Hello guys, what's up? So here I am again. We are going to do a complete CA foundation marathon. So this time people, it's not just going to be marathon. There is a lot more coming your way. Now in this video, you're going to find all these being covered. Now what is that when I say all this? 100% syllabus coverage, you can be rest assured. The next one is ABC analysis, which chapter is important and how many marks you can expect from each chapter. Even I've tried to cover that. The next one is people, very important people. I've tried to discuss all the case laws. When I say all, 100%, even just one line of a case is given in your CA Foundation ICAI material. I have discussed that. So I've discussed all the cases completely with facts. What was the provision and what is the conclusion of that particular case. I've discussed in detail and I'm telling you, don't miss this. Very, very important. And along with that, I've covered 5 RTPs, 5 MTPs. You can imagine, just sit back, relax. So those many questions are covered. And not only that, people, I've also covered some tricky questions which you guys may get confused, which is not seen anywhere but very, very important from your exam point of view. I've covered that. And not only that, the last part, I've also written the answer along with you, along with the student. I'll be writing and I'll be practicing that so that you guys will get a hands-on experience of how to present the law in your exam. So people, these are the things. Wherever possible, I will try to provide you the material. But remember, now the case law discussion and all of this, I will not be able to provide you the material part. So if it is not provided, please just don't ask the material part. So in this, I will not also be attaching the chart notes. It will not be provided. So the rest of it, please do ensure you just go through, enjoy the session, and wishing you guys the best throughout the session. So thank you so much and let's begin. Let's start your CA Foundation Law Marathon. Yeah, I don't know. We'll try to touch every topic. Wherever, again, in every place, every revision, I tell the same thing. If you guys think there is some topic which is very difficult, you can let me know. We'll try to go in detail in that topic instead of just as a revision. We'll try to go in detail for that particular topic. And this time, let us try to cover more questions also inside the class as and when the topic is done. As and when a unit is done, let us try to see some tricky questions that has been asked in the past. And you also will get a fair idea whether your mindset is properly working towards the question or not. And yes, let us try to do some ABC analysis. Which chapter is more important? Which chapter is less important? Let us try to do that as well. And I'll try to give you one sections chart, which is again important if you guys are planning to remember sections, because I don't know in which stage of your revision you guys are in. But I believe if you guys write 1 or 2 section numbers, because you all will have that question, right? Should we write section numbers in law? Correct? We have that particular question. First of all, how many of you are willing to write section numbers? How many of you are not willing to write? Meaning I'm not able to remember. Okay. Very hard word. Remember, when I asked you how many of them are willing to write, you saw the number of hands going up. Now, because they are writing, you should also write. Yeah. So either convince the entire country, don't write section numbers, or you start writing it along with them. Of course, I'm not saying at your level, if you write or if you do not write a section number, they will deduct a mark. I'm not saying that. But definitely a person putting that effort in writing a section number will definitely be given a little more weightage when compared to a person who is not writing section numbers. That difference will definitely be there. And don't you think it's fair enough? It should be there, right? A person who is putting the effort to remember the section should be given that 1 extra mark, right? So I'm not saying that you will lose a mark if you do not write a section, but a person who is writing a section number will definitely have that advantage. Now, is it possible for us to remember all the sections? Definitely no. So what we need to do?
Now, there will be so many topics which you guys would have come across saying that this is important. Now, whenever it is important, you make your note. Go towards the end. Write down that particular section number. Mark it in your book saying that it is important. Now, if you guys do it from your end, try to remember sections for that particular topics at least. Now, when they're asking that, you should be able to write. So, I'm not expecting you to write section numbers for whatever 24, 30 questions that is asked inside the exam. I'm not expecting that. But doing this, yes, it will have some extra advantage in your level of your exam. Yes, point number one. Point number two, people, fortunately or unfortunately, I don't know, law has been the most difficult question to crack for a lot of people. It is becoming a bottleneck. Law will be difficult. Now, why? Is law difficult or what is difficult? Remember, understanding of concepts is not difficult. You guys are understanding the concepts. Then where is the technical or where is the challenge coming? Remembering is there where the challenge coming? The answer is no. You guys are not getting an art of how to write. That is where the difference is happening. Why? Now, my question to you as we sit, how many questions have you guys practiced writing in law? How many? How many has not even opened one question yet? I've not practiced writing even one question. How many of you think I didn't even write one? You all have written quite a number of questions. Okay. Morning, morning, Panchayati. Panchanga and all came up. Now, okay. Yes. So, why I'm saying that is okay. I don't know how many questions you guys have written. You need not even have to tell me. But remember, people, the more you write, the better for you. Now, from today, have a task. At least write 3 questions in a day. At least three. Now, what do you want me to do with that three, sir? Remember, people, take a random question. Now, you do not even want someone to give you that. There are past papers, there are RTP papers, which is there right available in your book only, in your website only. Yeah, download that. Write down a question, write down the answer, and compare with the suggested answer right there. If you guys are trying to go somewhere nearby, well and good. If you are not able to go nearby, that's the challenge. And that's where we currently are. And that's the reality check. Yeah. And I'm telling you, the last time, though, the result was in law, it was very pathetic. Yeah. So, where the difference happening, it's there only. So, there are two differences, two ways. Remember, one, you give your attempt. After that, you realize, so this is where my mistake happened. And I'm telling you, this is where mistakes are happening. Try to correct it. Are you getting the point? Yes. Practice as much as possible. If you practice more, the chances of you scoring more is always there. Write down tests. And remember, the third challenge that you will come across law. For people who have given attempts, you will know. Time. You can't, I'm telling you, completing 100 marks is impossible. As a teacher, I'm telling you, there's a difference between something called difficult and impossible. Agreed? And I'm saying it is impossible. You can't write 100 marks. It is going to be lengthy. Now imagine when I'm already making that statement, you directly going to the exam on that day and writing your first paper directly in the exam hall. You remember and you try to imagine how the difficulty level will be. Hand won't go forward. The more tests you write, the better for you. The more you write, the better for you. Getting the point? These are all the mistakes that students do. And at the end of the day, you will feel no, that something went wrong. Nothing would have gone wrong. The planning is wrong. If you get all these right, it is not something which is very difficult or something. The third thing, now for example, uh, now they expect you to write one answer. Now in that answer, people, there will always be something called as a keyword, a provision, the main word. Now, for example, I'll ask you, what did you have for your breakfast? Now, the answer has to be idli, dosa, or whatever you guys had. Now, what will you guys write? Sir, I had, like this, the new restaurants. How do they define the dish? I had the rice batter added with lettuce, dal. Now, that is what you guys are writing. Dosa is the answer. But what you guys write, the most complicated way of presenting. You know how? I'll just try to run the words in my mind, in my own language. That I will just convert and translate into English. Hey, you evaluator, you do whatever you want. This is the answer. Exactly cut, copy, paste is a scenario. Now, is it a challenge? Yes. Agreed. I'm telling you. Now, there are three other subjects in your, foundation. Those three are not testing your language. This will test your language also, unfortunately. Now, should we do something for that? That's why I'm saying you writing practice will help. Agreed. So remember, I'm not scaring you, but people, this is how it is going to be. It will be difficult. And why? If I prepare you for a difficult attempt and if the attempt comes easy, then I'm the happiest person. But if I tell you people it will be easy, da yo go da chill, you will chill more. Huh? Let that not happen. Agreed. There was one student people who has got around 90 odd in QA and 90 odd in economics, 88 or something in what are that accounts, and 36 in law. I'm telling you, even if it was a 40, should have been a AR1. Yeah, I'm not scaring you. Sir, you are. That's why I'm telling you. That's the intention. Of course. Yeah. Why? Because for the next 12 hours or 16, I don't know what is the time, the way you look at the monitor should be different. It should not be with the chill, relaxed mode. If that is the case, I'm telling you the result now only. I don't want to prepare you. Macha, illada, ella okay. Always welcomes you. That and all I don't want to do. No wrong setting of the trend. This is the trend. Yeah. Now accordingly you prepare. You have time. You have ample amount of time. Don't think that I've wasted so much of time till now. All that is okay. Done and dusted. What is there in your hand? Try to focus on that part. Are you getting all of you? Yes. So try to focus on that part, and yes, the rest and all will definitely be good. Yes. Okay. So am I audible online? Online. Everything is good? Okay, perfect. So the first thing most of you will have is what is the weightage? What is the weightage? Sir, first thing, which one should I skip? You tell us which chapter we can skip, then write off that chapter first. Now I'll tell you what is the weightage. You guys plan it accordingly. Now this is how your uh, index look. Indian regulatory framework, one question, 6 marks, pakka. Huh. Yes, now. Now we will see. Indian regulatory framework, you can expect around 6 marks to come from Indian regulatory framework. That's the weightage of the first chapter. One question will definitely be there, and at least in the last 4 attempts, it has been proven that it is going to be a direct question. They will directly ask you what is the source of law. They will directly ask you what is the Supreme Court, High Court. It will be a direct question. So do not skip this. The most easiest one to tackle is this particular question. Do not leave it. Now, next coming to your Indian Contract Act, you can expect somewhere between 30 to 32 marks. That is your Indian Contract Act. 30 to 32 marks. That's the weightage. So never skip anything in Indian Contract Act. Now, Sale of Goods Act will come to around 22 to 24 marks. That's the higher limit. The Sale of Goods Act will come around 24 marks. The next one is your Indian partnership. You can expect anywhere between 18 to 20 marks. That's the weightage of your Indian Partnership Act. LLP Act, again, there will be one question for sure. It will be somewhere around 6 marks. Companies Act, anywhere between 20 to 22. Let us write, say, 21 marks. Negotiable Instruments Act, there will be somewhere around 14 marks. Yeah. Or you can write, say, 10 to 14. Yes. Maximum, minimum, comparing everything, that's the weightage. Is clear? Yes. Now, sir, which one can we leave? Don't leave anything. But no, sir, please tell us. I will not tell what to leave. I'll tell you what is more easier to concentrate. Indian regulatory framework, easy, direct question now. Hardly if you guys rattamar, meaning literally memorize. Even if you guys are able to do it for say 8 pages, that's the volume of the chapter. You will pakka get 6 marks. And very assured, do not leave this. The next chapter you should never leave. Which one? LLP. Don't leave a cakewalk. There will be there is nothing there to test. Some 6 papers, 7 pages, if you read and go, pakka you will get 6 marks. Don't leave that. I'm saying in these chapters, you need to get out of out. If they're asking one question, 4, you need to get 4 on 4. If they're asking it for 5, you need to get 5 on 5. I get in the point. Yes. And the next one, what is the next important one? Which one? Yes, sir. Very good. Companies Act. There is no practical aspect at all. Questions are more predictable. Now, where are you guys getting confused? Indian Contract Act. Sir, we don't know which provision only. Then what is the easier one? Companies Act. Agreed? No. I don't know if you guys have gone through Companies Act. If you ask me, yes, that's the easiest one of all of this. There is no confusion between whether is it Indian Contract Act or Sale of Goods Act. Now, in Indian Contract Act, we will get confused, sir, which provision. Nothing is there. No headache. Now, people, if you guys do this only, if you do this properly, then you are almost getting 35 marks. Now, what is that you need to handle? Now, you tell Indian partnership, is it difficult? At least 2 direct questions will pakka be there. Now, out of what? What is the Indian partnership? 18 to 20. At least 10 to 12 marks direct question will be there. Now, 35 plus 10, how much? 45. I have not even touched no Indian Contract Act till now. Now, out of Indian Contract Act and Sale of Goods Act, which is having a weightage of around 55 marks, can't you guys score some 20 marks? 55. For every 5-mark question, can't we score 3 marks? That's all, no? You will get exemption only, no? Sir, theoretically everything will be correct. Practically, bunny exam, you will know. Huh? Yes or no? But why I'm telling you is try to concentrate in this order. It will help you. When you're seeing this particular question also, you should not go wrong. Getting the point? Hello. This is your ABC analysis. If it is going to help, then go ahead. This is how it will work. Clear? Okay. So agenda for the day. Let us do Indian regulatory. Okay, well, let us do whatever we can do. Let us do it, and we'll try to solve some questions also. Then we'll see. Yes, all of you. Okay. Let us start with the first chapter, chapter 1, Indian Regulatory Framework. Now, what is the Indian Regulatory Framework? Online, is it okay now? Online? Is it audible now? Fair enough? Okay. Okay, perfect. Okay. Now, people, Indian regulatory framework. Now, what is there in Indian regulatory framework? So, technically, there are 3 people regarding whom you guys will be studying. We also call them as Three organs of our government. Now, what are the three organs of our government? There are three things. What? First one is called legislature, executive, judiciary. What is the role of legislature? Legislature's role is what? To make law. That is the first question. Two times they have asked. What? What is the source of law? Or what is the process of making law? Two times they have asked. Direct question, 6 marks. Simple, huh? There is nothing, no invention, no nothing to be done. Directly they'll ask her. No usage of any practical, nothing will be required. Getting the point? That's how direct it will be. Agreed? Okay. Now, okay, let us start. The three organs of government, one is called as legislature, one is called executive, one is called as judiciary. So there are three organs of this government. Now, the first one is called as legislature. What is legislature? Legislature is nothing but that is where the law is made. This is nothing but people, parliament in the central level, in the state level, we call it as state legislature. You guys call no Vidhan Sauda, Vidhan Parishad and all. That is where the law is made for states. For center, where is the law made? The center, the law is made in parliament. What do you mean by parliament? Lok Sabha, Rajya Sabha. Now, how do they make a law? To make a law, what do? They first think that, let us imagine, not everyone will know every subject. If you ask me what is my knowledge on QA, I'm not sure. I might even very well fail also. Yeah. Now, but what if it is law? That's my strength. Like that, don't you think for every subject matter, there are people who will have that as their strength? Now, what we will do, first the government will identify where do we need to make a law. And they will identify a person and they will call these people as committees. They will form a committee. Now, this committee, him along with another 2-3 people, they will make all research possible and they will give something called as the first draft. Meaning they will give the basic version. Now, this basic version will be first introduced in Lok Sabha. All our ministers sitting there, they will debate on it. They will eliminate points which are not required. They will come up with suggestions. All those suggestions will be inculcated. It will be taken, inside. They will change. They will modify. After they approve, okay, now it is good. It will go to the next house. That next house is called as Rajya Sabha. Again, they will debate. Again, there will be a debate. Again, people will take time. Again, modifications will happen. And finally, they will give an approval. That is how Rajya Sabha approval will come. So once it is agreed, the draft is agreed, or we will also call it as a bill. Once the draft is agreed or the bill is agreed, now it will go to Lok Sabha, Rajya Sabha. After both of them agree people, it will now go to the next person. That person is called as President of India. The President of India will now look at that entire draft that Lok Sabha, Rajya Sabha has approved. And what will President of India do? The President of India will sign this particular bill. Now, it is all in the center. We don't know what is happening. How will we all know that this law is implemented? They will put it in one book. That book is called as people Official Gazette. Official Gazette is nothing like a newspaper. Da. If it is coming there, then it's a message for the entire country that this law is implemented from today. So once any official gazette notification comes from that day, that means that law is official. From that day, the law takes birth. Now, this is what is called as what? The process of making law. This is what is the question they have asked. So what is the process? First, it will be a committee will be formed. A committee will come up with a draft bill. The draft bill will be introduced in Lok Sabha, that is both houses of parliament. Once Lok Sabha gives its approval, next it will go to Rajya Sabha. Once Rajya Sabha also gives its approval, it will go to President of India. After its approval, then it will go to Official Gazette notification. That's the process of making law. Yes, sir. Specialized committee is formed to draft a bill on the subject matter. The bill shall be presented in both the houses of parliament, Lok Sabha, Rajya Sabha. Such will be now given to President of India, Official Gazette of India. Is this clear? Now, what is this union list, state list, and concurrent list? Heard of it? Nothing but people who should make law on which matter. Now, for example, there is something called as uh, GST. Who should make law? Is it center? Is it state? Who should make law? For example, education. There is agriculture, or so many matters are there. Who will make a law on all these matters? So, to avoid confusion, in Constitution of India only, it is clearly written, people, who has power to make law on which subject matter. They have written clearly, okay, list A. If at all a particular topic is coming in list A, then only the center has a power to make a law on it. Now they have written something called list B. In list B, if a topic is coming, only a state can make a law on it. Center will not make a law. The third list, if at all a topic is given in third list, then people, center and state, both has a power to make a law on it. Example, if it is finance, Feb, budget, it is only with Nirmala Sitharaman. Will Sidramaya speak on it? No, because it is central. It is center, and that's why everything is going in union list. State list, agriculture. That's why if you go towards, nowadays it is less, but 5 years, 10 years back, farmers would have taken loans. Whenever new government comes, they will say, we are waiving off all the loans. Center is not having that power. It is your state specific power that is there. If you want, you will decide. The third one is concurrent, education. You have no state syllabus, central syllabus. Both has power to make a law. So accordingly, the law will be made. If it is union list people, the law will be made in parliament. If it is state list people, the law will be made in state legislature. That is what is called as your Vidhan Sabha, Vidhan Parishad, Vidhan Saudha, whatever you guys know. That is only called as state legislature. The third thing is called as concurrent list, where both of them can make a law. Is this clear, all of you? Hello? All of you? Okay. The next one is called as people types of law. There are almost 4 types of law. Now, what is that? First one is called as criminal law. Now, what do you mean by criminal law? Criminal law is nothing but people. What is criminal law? Huh? What is criminal law? What is criminal law? Criminal law is, see, there are generally people, 2 wrongs that can happen. There are 2 wrongs. One is called as public wrong, one is called as private wrong. If at all any public wrong is happening, we call that particular act as people's criminal wrong. Now, what do you mean by that? For example, let us imagine yesterday 8 o'clock, one person was walking on the road right in front of our academy. Now, someone came and killed that person in the most brutal way possible. Now, you tell me, after this incident, for the next 1 month, no one will walk in this road at 8 o'clock going forward. Agreed? Yes. Now, people, this is called as what people public wrong. Now, why? See, someone has killed someone. Yes, that person passed away. But that impact will be there on the society. Society will lose, what is that? The faith they have on the system. They will start doubting the police. What are you guys doing? We will lose faith over the system. And that's why, remember, if it's a criminal wrong, who will fight your case? You will not fight your case. The person who passed away, he will not fight. Of course, he will not fight. His family will not fight. Then who will fight? The government, the state will fight your case. That's why people, all the cases, now for example, Darshan's case, it is state of Karnataka versus Darshan and others. Yeah, Delhi case, Nirbhaya case, it is state of Delhi versus Mukesh and others. Why is Delhi fighting? Why not the family? In criminal law, remember, injustice happened because of lack of control over the government. The who has failed in their job? The government would have failed. The police would have failed. So they will fight the case for you. You will not fight your case. That's how the criminal law works. Yeah. Now imagine this person was killed yesterday. We will give him some his family. The person whoever killed, he will come and say, Anyways, the person is gone. I will give you 50 lakh rupees. Settle the matter. Don't go to court. Is it okay? Why? Imagine even in court, I will go and say, sir, person is gone. Now, for example, you know the famous murder that has happened, the celebrities murder and all, whatever has happened. Now, let us imagine if someone comes and says, we will give compensation. We have money. We will give 1 crore as compensation. Okay, can we settle it? Why? Now, money, see, anyways, the soul will not come back. The person has passed away. That person will not come back. So, can I give money and settle the matter? Why? We can settle the matter, no? Criminal cases can never be settled. Now, why do we go to court in the case of murder, in the case of theft, in the case of kidnap, rape, whatever is the scenario? Why do we go to court? We go for justice, not for compensation. There is difference. You go for justice. Now, what do you mean by justice? Justice is, sir, this person was affected, punished. I want even this person also to be affected and punished in the same way. So you guys go to court for revenge, not for compensation. Criminal case, what you ask in return is jail, capital punishment, hang him. Hello, understanding? Now let us imagine you guys go and eat some food on in some hotel. When you guys are eating some food in hotel, let us imagine people in that food, there is some foreign object. Foreign object, sir. Foreign means someone, foreigner is there. Foreign object, let us imagine some bee is there, some insect is there. What will you do? Appapa, latre. You'll be happy? No? Now, people, what are you saying? You're going to court, you're filing a case on the person, and you're saying, sir, do one thing, hang that chef. Hang him, sir. You tell me, is it right? Why? Why, da? Hey, you should be thankful, da. You got one extra object, Huh? Along with one potato, onion, you're getting one B. Then who will give you? He's concerned on your health. Yes or no? Now you tell me, what will you go and ask in the court? Sir, take this vada, give me one more vada, that's all. Huh? That's what you want to know. Remember, people, this is called civil case. Civil case, what you guys need is not justice. You guys need compensation. Macha, your chapter, breach of contract and its remedies, was there hanging there? Capital punishment, put him in jail for 20 years. Was it there? No. Then what was there? Ordinary damage, special damage, exemplary damage, vindictive, nominal. Why that? Because what you want is money. End of the day, whatever is the name given, in all these, you are getting money only in return. This is the difference between criminal law and civil law. Understood, all of you? Got some fair idea? Hello. Criminal law, you always want justice. Who will fight? You will not fight your case. The state will fight your case. And what you will get in return is capital punishments. You will get imprisonments. Whereas in civil, what do you get? You guys will get compensation, money. These are called as civil cases or civil law. These are called as criminal cases or criminal law. Now, in India, what are the criminal laws? Which one governs the, what is that? Laws. Your, you guys can write this also. IPC and CRPC is replaced also. I hope you guys know. So I think in IPC and CRPC, we used to write this. You can have it in your book, make it a point. Somewhere you write it because it is implemented as well. Yeah. So we had two laws which used to govern our civil and criminal cases. I mean, specifically, I'm saying criminal cases. And that was called as IPC and CRPC. Today, IPC is replaced by BNS, Bharatiya Nyaya Sanhita. And CRPC is replaced by BNSS, Bharatiya Nagarik Suraksha Sannita. Yes, sir. So earlier we had two laws, IPC, CRPC. Today it is replaced by these two things, BNS and BNSS. Clear? Copied all of you? Done? Okay. So that is what is given here. Criminal law, it is a law relating to violation of public wrongs. It is governed by BNS, BNSS, which defines with crime, nature, punishments under IPC and procedures for executing the punishment under CRPC. So what in BNS it says, if you guys do murder, then the punishment will be say imprisonment for 14 years. BNSS says how should this trial happen? Within how many days you have to bring him to the court? Within how many days he should be arrested? Evidence has to be collected. How the procedure is given in BNSS. That's the difference. Okay. Next one is civil law. Law related to the matters of disputes between individuals or organizations. It focuses on dispute resolution rather than punishment comes under criminal law. Administration of civil law is by CPC. It can be classified into law of contracts, family law, property law, and torts, etc. So breach of contract, everything will come here. Murder and everything will come under criminal law. Clear? Next one is called as common law. What do you mean by common law? Common law is nothing but people. What is Balfour versus Balfour? Carlyle versus Carbolic. Raman Shukla, what is that? Lalman Shukla versus Gauri Dutt. Your Salomon versus Salomon. What are all this? Case laws. Now, why are we learning these case laws? What is the use of it?
Because judgment can be given to the similar cases.
Okay, so whenever imagine people, you have already seen, if at all someone is killing someone in this way, then the punishment earlier was 14 years. After some 5 years, someone again kills one more person in the same way. Now, I need not have to reinvent the wheel. Already in one case, they have already clearly given, if you kill someone in this way, then the punishment you will get is 14 years. Let us imagine 6 months back, there was one hotel where I told you the incident. It is a real incident that a person was, he ordered for some Bisibelabath. He got an object in that particular Bisibelabath. That person got a compensation of 65,000 rupees. Now, what will I do? Now, imagine you guys go in the break. You guys have a breakfast. In your breakfast also, the same B comes. Yes, sir. Now, there is already a precedent. Sir, 6 months back, in one of the case, same incident happened, and that court, they gave a judgment that you will be entitled for 65,000 rupees as compensation. Can I also get the same thing? The judge also will say, because the facts are same, I will give you the same particular judgment, and hence you will also get same 65,000 rupees. Now remember people, whenever in the exam, you guys would have studied so many cases. If the story is similar, you are expected to write the name of the case. Sir, is it optional, mandatory? It is mandatory. But the story has to be same. What do you mean by that, sir? So in that case, it was Bisibelabath. Here, my case, it is Dose. His story is same. They same only, da. Food is changing, that's all. Story is same only. But sir, that was Bisibelabath. This was murder. Can I put the same case here? No. Same thing will apply to your exam also. If the case is same, you are expected to write the name of the case. If it is not, don't write. Is it? You're getting the point?
Yes, sir.
Writing the case law name will definitely give you an additional mark. It will have weightage. Are you getting the point? All of you? Now, for example, if there is a question on domestic agreements, husband and wife, close your eyes and write off Balfour versus Balfour. General offer, open offer, right of Carlyle versus Carbolic Smoke Ball Company, minor, right Mohri BP versus Dharmodas Ghosh. That's how you need to think. Getting the point? Hello? Okay. Now, common law is people that, what is this? It is called as a judicial precedent. That means what people? Case law, which is already decided by the court, is called as people common law. There is one article in Constitution of India. That article is called as section one, Article 141. What do you mean by that Article 141? In Article 141 of Constitution of India, it is clearly written, people, that if Supreme Court decides anything, it will bind, the same decision will bind in the high courts, in the district courts, whatever the lower courts, they will have to follow the decision given in the Supreme Court. And that is what is called as common law. Hello? Are you guys understanding? So if Balfour versus Balfour, they have clearly given any contract between husband and wife, it is clearly given as domestic agreement. Tomorrow, if any scenario, similar case happens, we go to the court. You can give Balfour versus Balfour as a judicial precedent. The same judgment will be given in your judgment also. Getting the point, all of you? Yes. Okay. Next one is called as, in common law only, they have given the word called as stare decisis. What do you mean by stare decisis? Yes, Divya, you have to write that BNS. Write that BNS. Stare decisis means people nothing but to stand by what is already decided. So if it is already given, one court has given a judgment, whatever has been given there, same thing will apply here also. Cut, copy, paste, nothing will change. Clear? Yes, sir. Okay, done. Next one is called as people principles of natural justice. What is my principle of natural justice, people? Two things are important. What? It is given in our movies also, no? What is that? You should not be a judge of your own. A comes and kills B. Now B's brother will go and kill A. Is it fine? Answer is no. That is what is the meaning of don't become a judge of your own. You should not do what is right. You have to come to the system. System will do what is right. Now, sir, there is an allegation that A has killed B. Can I directly pass an order? Go and hang A. No. You have to call A to the court. You have to give an opportunity of being heard. The best example I can give you is the recent murder case going on. So many evidences, so many things. But are we passing an order saying that, yes, you are the culprit? Are we passing? No. That's the exact meaning of audi alteram partem. What is audi alteram partem? Audi alteram partem is nothing but people opportunity of being heard. A killed B. Now I should ask A, why did you kill B? I should ask why? Because what if it was a self-defense? So many questions will come. That's the simple thing of something called as audi alteram partem, and that is only called as common law. Common law is nothing but people. I have to give the opportunity of being heard to the culprit before I pass any order against him. That's the basic common law. It is also called as principle of natural justice. I cannot pass an order arbitrarily. I cannot just say that, yes, you will be punishable under law. Yes, you only did the murder. You might have done it, but I have to give you an opportunity of being heard. That is only called as common law. Understood, all of you? Tell me what are the four laws. What is the first law? Criminal law. What is criminal law? It is anything which is public wrong. Write down those points. That is what I call as keyword. Now I asked you criminal law. Now you know what is criminal law, but you are not able to write the points. You're getting what I'm saying? Now you know criminal law. Write down the points then. First one is public wrong. Second one is what you seek is punishment, not compensation. Third one, who fights your case? State fights the case and not the individuals. And the fourth one, it is governed by the law. BNS, BNSS. What is civil law? It is a private wrong. It's a dispute between individuals or individuals and organizations. Okay, what is the remedy you want here? Compensation, money, and not punishment. And yes, CPC is governed here. Okay, and what is the third law? Common law. What is the common law? What is the word you will use? Stare decisis. Meaning what? To stand by what is already decided. And it is also called judicial precedents. Okay, the last one is called as what? Principles of natural justice. Audi altrum partum. Meaning what? Giving an opportunity of being heard. Hello? Yes? Are we good? Yes? Okay. The next one is called as people executive. Remember, people in executive, there will be a question. Pakka. There will be a question in executive. What is executive does? Enforcing of law happens by executive. The best example I can give you is people police. Now there is a law that you guys have to wear helmet. You guys have to do triple driving. Correct? No. He's saying, yeah, 4 people, sir. What triple? Triple and all done long back. Now we do 4 only. There is at times I wonder, is there a difference between share auto and the boys ka bike? Share auto will be taking less people. Boys, macha ba, silencer, there is still some space. Hold it. Huh? Friend, sit down, macha. You only. I'll put one seat for you. Noda, boys. Yes, sir, noda. The circus acts irutte. One person will be there. Ingon kite kondu, that person will be hanging. This person will be hanging. All these things you guys will do. Now, people, that is what they are telling you what. Now, whenever there is a law, don't do triple driving. Don't do, what is the driving without helmet. Without DL, you cannot drive. All these laws are there. Will you guys follow? Will you guys follow? Will you follow? Ayo, sir, depends, sir. Ali, police mama, police, police inspector, if they are there, then you will follow. Yes or no? See, this is road. Illi, the police uncle will stand. People, they are standing people for our own security, safety. But see how unfortunate our country is. If at all they are standing there, we act like magnets, repel. Wherever the police uncle stands, there will be automatic deviation of vehicles. We will not go there only. Why? I don't know. Correct, Noda? Yes or no? Beauty of the country. Okay. Now, what is this person doing? This person is called as enforcer of law. Because he is there, you're going with law. If not, will you go with law? Na? Illa. Iyo. Correct? No, share ata only. That's what is called as people executive, the one who implements the law. Example. Now, SEBI, you have to follow SEBI laws. If you're a listed company, but will you follow? Answer is no. So what did we do? We formed a body called as SEBI. SEBI implements the law. If you guys do not follow the law, SEBI will give you punishments. So that is what is called as what people? Executive. Executive's role is what? Law is there, but it will make sure that the citizens will abide by the law. How? At times with words. If not, at times with lati. COVID, don't step out. Did you guys listen? No. One tapak, then everyone listened. So that is what is called as what? Executive. Executive will always implement the law. They will make sure you are abiding by the law. Agreed? All of you? That's the second role, the role of executive. There are too many people that has given here. They'll directly pick one question. They say, for example, they will say Ministry of Finance. They will ask a question. What is the role of Ministry of Finance? They will ask you a question. What is the role of Ministry of Corporate Affairs? Directly, you can expect a question. Yes, remember and go. Important. Enforcing, executive only, you can expect one question. Important. No and go. Yes. What is Ministry of Finance done? Vitta Mantralaya. What is Ministry of Finance? They take care of your finance. Your budget, whatever your transactions, see, end of the day, there has to be someone who takes care of expenditure of the government. Now, in our home, our mother or father is taking care of it. Now, they are the in charge of Ministry of Finance. Same way in India, we have something called as Department of Earning, Department of Spending. Who will overlook these two departments? It is Ministry of Finance. Those departments only is called as Department of Earning is called Department of Revenue. Department of Spending is called as Department of Expenditure. Now they will take care of everything. Now government has extra money. What to do with extra money? Department of Investment and Public Asset Management. Now this month we have extra money. Next month we might need money. Now you guys will invest in savings bank. Who will do it for government? It will be done by the Ministry of Finance. That is their role. Next one is what? Department of Public Enterprises, meaning whatever the public enterprises are, the expenses of those public enterprises, the operational aspects, they need money to run. Again, it will be taken care by Ministry of Finance, Department of Financial Services, Department of Economic Affairs. All these things, anything to do with money, it will come under Ministry of Finance. Next one is what? Ministry of Corporate Affairs. What does MCA do? There are some acts in India. One is called as Companies Act. One is called as LLP Act. One is called as IBC Act. Companies Act, LLP Act, Insolvency and Bankruptcy Code. Now, Companies Act is there. What is the guarantee that they are all following all the sections of Companies Act? What is the guarantee? What they do is, see, on the top people who sit, the person who sits in the top is called as central government. Now, central government means what? What do you guys think of central government? One person that comes to your mind is Narendra Modi. Can Narendra Modi do everything? Department of Education, Department of Tourism, or Department of Culture, can he do everything? No. Now, what do? We try to segregate the duties, and that is only called as what people departments, or you can also call it as ministries. For example, finance. Narendra Modi need not have to take any decision. Why? We have appointed a specific minister for finance, and that person only is called as who? Nirmala Sitharaman. Now, Narendra Modi won't come and do anything there. That department, that ministry is given to her. In the same way, in India, Companies Act or corporate matters, again, Modi need not come and take a decision. We have formed a ministry for the corporate, body corporates, and that ministry is called MCA, Ministry of Corporate Affairs. Remember, same minister is the minister of MCA also. Nirmala Sitharaman is the minister of MCA as well. Hello? Now, any decision with regards to Companies Act. Now, for example, what do you mean by a small company? What is a small company? Paid up capital not exceeding 40 crore. Turnover not exceeding 400 crores. That's small company, big company, 400 crores and all you guys are giving limits. Paid up capital is 4 crore and turnover is 40 crore. Is it and or? Or any one condition to be satisfied? And or? Pakkana? Exactly 4 crore, exactly 40 crore. Is it a small company? Paid up capital is 4 crore. Turnover is 40 crore. That's the answer. Correct. Exactly a company has 4 crore capital, 40 crore turnover. Is it a small company? Okay, how many of you think yes, it is a small company? Exactly 4 crore, exactly 40 crore. How many of you think it is not a small company? Exactly 4 crore, exactly 40 crore. It's not a small company. Exactly 440. Remember and go. What you remember and go is at 440. The question will not be 4 and 40. Questions will be around the words. What is a small company? And you will forget. Is it and or? Both conditions to be satisfied or any one condition to be satisfied? That you will forget. Yes or no? That's where the mistake will happen. It's and, not or. Both conditions are to be satisfied. Paid up capital not exceeding 4 crore. So up to 4, you're a small company only. Turnover not exceeding 40 crore. Up to 40, you're a small company only. But remember, today's small company means 4 and 40. What was small company 2 years back? Huh? 50 lakhs? So people, this limit did not become 4 and 40 immediately. It was 2, 20, 50 lakh was there. Now everything, it has changed with time. Now who made this change? Now that is where people, we need someone, no, MCA will come and make the change. Hey, today life is changing, da. 1 crore is no longer small. They said 2 crore. Hey, 2 crore is no longer small, da. 4 crore. I'm telling you, next 2 years, it will again increase. Who will make this change? Central government. That is the role of MCA. Understood? What is the role of? Hello. Executive implementing the law. Understood? Hello. Okay, next one. Ministry of Home Affairs. What do? Ministry of Home Affairs. What do? Jihad, terrorist, discount. Correct? Your nation's safety, security, all your internal securities, everything will come under them. See, remember, Griha Mantralaya, departments of Ministry of Affairs, what and all will come under them. Easy to remember. What and all is easy to remember. Border management, easy, Internal security, easy, When I say border, one person will by default come. Easy, So easy to manage, Yes, sir. Next one, Home Minister, Home Affairs. So Department of Home will be taken care by them only. Next one is Department of Official Languages and Department of States. So these are the departments that come under Ministry of Home Affairs. Remember and go. Next one is called as Ministry of Law and Justice. Now, what is Ministry of Law and Justice? Imagine people, someone files a case on the government only. There should be some policies, process to take or defend the governments. Who will defend them? Their lawyer is called as people Ministry of Law and Justice. What will they take care of? They have three departments. One is called as Legislative Department. Next one is Department of Legal Affairs, Department of Justice, respectively. They take care of any cases filed against the government and every administration around that. That will be their role. Next person is called as SEBI. I need not even tell you what is SEBI. Anything with regards to stock market. We have appointed one inspector to check everything with regards to stock market. That is this person's role. Agreed? Implementing of anything regarding stock market. This person is called as SEBI. Listing, IPOs, FPOs, stock exchanges, insider trading, Satyam scam. And what is that? Scam 1992. Arshad Mehta. Everything will come under SEBI only. Because of that person only, this person took birth. Arshad Mehta, Anna, see how powerful. Next one is RBI. Whatever is the eyes here for stock market, same eyes, cut copy paste will be for simple, Simple. That is only the role of RBI. See, same thing I'm explaining you. In every place, what is the role they are playing? They are playing the role of a cop. For us, the traffic police was a cop. For the banks, RBI is a cop. For stock exchanges, SEBI is a cop. Because SEBI is there, these people are implementing the law. They're following the law. Banks are following because RBI is there. I think that's why they are called as executives. Hello? It's a central bank and regulatory body responsible for regulation of Indian banking system. It is under the ownership of Ministry of Finance only. It will come under Ministry of Finance only, RBI also. It is responsible for the control, issue and maintaining, supplying of Indian rupees. Remember, chances of RBI will be more. You guys want money in circulation. Who will control that? Comes under RBI. Printing, Mudrana, comes under RBI. Notes, someone has to print, no? Open notes, it will be there. Reserve Bank of India. Yes or no? It also manages the country's main payment system and works to promote its economic development. Now, if you have to make a payment, you will tell your bank that I'm scanning for a tea. 15 rupees has to be made. Your bank will make the payment to the 15 rupees. Agreed? For government, who will make the payment? RBI, government accounts will be with RBI. Any money to be received, it will be taken care by RBI. Hello? Bharatiya Reserve Bank Note Mudran is a specialized division of RBI through which it prints and mints Indian currency notes. Print is for notes, mints is for coins. And two of its currency printing press located in Nashik and Devas. Coin, again, there is a little, different departments are there, but for us, this imagine it is coming under RBI. RBI established National Payment Corporation of India as one of its specialized division to regulate payment and settlement system of in India. There's nothing but your UPI. You get the national payment system cycle. But yes, next one is Deposit Insurance and Credit Guarantee Corporation. What is this DICGC? What do they do? Now you guys have done your FD in one bank. Imagine you have done a FD in Axis Bank. What will you do if this bank fails? What will happen to your FD? Gone, huh? You have done FD, no? What if you have done an FD in Axis Bank and that bank shuts down its business? What will you do? That is only the role of what you guys are saying is called as insurance. Now RBI has formed one subsidiary company, and that is only called as Deposit Insurance and Credit Guarantee Corporation. What is their role? Axis Bank will have to take one insurance policy for your FD account. If Axis Bank fails tomorrow, this company will come and give you the insurance amount for your FD. Sir, how much I will get? The maximum limit is people 5 lakh. Of course, these limits are being increased. Now, who is doing this insurance? That is done by DICGC. That's their role. Whatever FDs, savings bank, whatever accounts you guys have in bank, it is secured up to 5 lakh rupees. That's why you all have to diversify. If you have 10 lakhs, don't keep it in one bank. So if I have 10 lakhs in the account, you will get maximum 5 lakh only as insurance, not 10 lakh. But what if I keep it in two banks? You guys can get back 5 lakh from each bank. Understood? Okay. Next one is IBBI. What is Insolvency and Bankruptcy Board of India? Okay, there is something called as people Insolvency and Bankruptcy Code, IBC, which is taken care by MCA. This is the Act, IBC Act 2016. Why do we have this? There was a person called as Vijay Mallya. He ran one company called as Kingfisher. Kingfisher had to pay money to so many creditors and banks. Now they did not get 1 rupee also. They all started crying. See? They all started crying. Now where should they go and cry? You tell me. On road? On street? Police station? Where? They do not have a designated place to cry. One person though, he wanted to go and kill only. Directly kill only. Now where do I go and kill her? Where? Somewhere I should go and kill, no? Now I have to put out my anger somewhere. Where? There was no place. That's why in India, liquidations was absolutely not governed. So for that, they formed one act called as IBC Act 2016. That's the name. Insolvency and Bankruptcy Code. You want to go and kill, you have so much of anger, go and tell them. You want to go and cry there. Whatever you want, go and do there. So a specific body was created. That's the act. Now, who will take care of this act? We need eyes. No, this is the act end of the day. The eyes, again, is called as Insolvency and Bankruptcy Board of India. Hello?
Yes, sir.
Understood all of you? That's the role of IBBA. And they work under MCA only. Clear all of you? Make sense? I hope you understood what are the executives. Remember, IBBA also, they can ask you a question important. No and go. Clear all of you? The same thing is given there also. So if there is any insolvency matters of LLPs, companies, individuals, It will be handled by this IBBI, insolvency matters. What do you mean by insolvency? So I have taken debt, I have not repaid. Those matters will be taken up by this board. That's what they would have written. Correct? Huh? Makes sense? Huh? So if Kingfisher has to make payment to the bank, they have not paid, the banks will go and file a case in IBBI. IBBI will give you a certain time to repay. If you don't repay people, the company's existence will come to an end. It will be bound up. That is how strict this board is. Understood? Yes. Okay. And the last person is called as people judiciary. Now, what does judiciary do? The structure of Indian judicial system, they have asked twice. What is the role? What is the functions of judicial system? What is the function of judicial system? Judiciary is nothing but people. The third organ. What is the third organ? Court. Correct? Judiciary is what? Nothing but court. So the functions of the judicial system, what do they do? First one, regulation of interpretation of act and courts. Meaning what, people? Whenever the police is telling that, sir, this fellow had parked his bike in no parking. Now the police has arrested you. Now he will file a case on you. You guys both will go to the court. Now what will the judge do there? He will say under what ground you arrested or under what ground you took this particular bike under your possession. I will say, sir, as per section so and so of Motors Act or Transportation Act. So I will clearly define. Now what will the judge do? The judge will read the law and he will say, yes, what you did is right, what you did is wrong. That's the role. Interpretation of act means what? Reading and implying, understanding the act. That is the role of judiciary. Second role, what? There is a fight between two people. Of course, the court will come and resolve the dispute. Third one is promote fairness amongst the citizens. Because they are there, you guys will not fight. Agreed? The next one under them is called types of courts. The first type of court is called as people. Go from here to there. First one is called as metropolitan courts. What is metropolitan courts? If at all you are a metropolitan cities people with a population of 10 lakh or more, then for your cities, there will be specific courts designed. So if you have any problem, imagine people, your school days, you had some problem. In your school, there was a class teacher, there was a HOD, there was, I don't know, principal. So if you have any problem, do you directly go to the principal? Don't you think there is a hierarchy? Same thing applies in the court also. If you guys have any problem, you cannot directly run to Supreme Court or High Court. You have to follow a hierarchy. You have to first go to the lowest court in that particular city and next to the highest court of the country. Not directly you can go. Hello? So what is the first court I can go? Your class teacher. Who is the first court? If at all you are from metropolitan cities, the first court you guys will come across is called as metropolitan courts. They are established in metropolitan cities in consultation with High Court. So now Bangalore has metropolitan courts. Now if I go to say Tumkur, they do not have metropolitan courts. It is one of the city districts. It is not there. So it is there in Bangalore, you will go here. If it is not there, what to do? Then comes the next court, people. The next court is called as district court. Hello? Now district court can be again, people, further classified. There is something called as, it comes below High Court. It deals with civil law matters. There is one more thing called as, people, court of session. This is for criminal matters. Now people, see here. What has happened to you? Imagine there is a now I want to file a case. The case can be of two types. One is called as criminal case. One is called as civil case. If it is criminal case, people, I will go to something called as court of session. If it is civil case, civil courts, people, I mean civil cases, I will directly go to district court. Are you guys understanding this? Hello? Yes. So First court, your class teacher people, in the case of criminal cases is called as court of session. In the case of civil people is called as district court. That's your class teacher. Now your class teacher says what you did is wrong. But you think, no, what I did is not wrong. The class teacher is wrong. For example, you guys will be playing cricket. The umpire on the field will say you're out. But the batsman says, no, I'm not out. Umpire is saying, Arey, this is my job done. I've been appointed to see everything and I'm saying you're out. You're saying, no, I'm not out. What will you do? You will go for that DRS in the court system is called as people appeal. So if at all you're not happy with what your class teacher said, you're going to your HOD. This process of appeal is there. No, same thing will apply even in judiciary. If you're not happy with what has been given by district court, you will go to the next court. That is called as people high court, the highest court of the state. Hello? Sir, I'm not happy with what even High Court said. What do I do? Finally, again you will go. Sir, again appeal. The last place you will go to is called as Supreme Court. Is this clear, all of you? Yes? Sir, even this I'm not happy. Die. Yeah? So, only up to one extent you can go. You can't keep going. I'm not happy. You should be happy somewhere. If three people are saying you're wrong then. The highest possible place is called as Supreme Court. Of course, there is only one place where there is an excuse. Even if Supreme Court says you're wrong, you can still go to a higher place, only in one case. But it will not happen everywhere. Not required for us, so ignore. Yes, sir. So, this is called as what people? Appeal process. Clear? Sir, so I cannot go to Supreme Court directly. Can I not go? Can I not go to High Court directly? Generally, no. You can't directly go to Supreme Court or High Court, but in only one case you can go, and that is people. If your fundamental rights are breached, only for that you can go to Supreme Court directly, or you can go to High Court directly. Only for these two. Sir, what do you mean by that? You have a right to speak. You have right to movement. That's a fundamental right. Now, if someone is taking away that right from you, you can directly go and file a case in High Court. You can directly go and file a case in Supreme Court. You need not have to go to District Court and all that route. Hello? Getting the point? Yes. So this is called as Supreme Court. This is called as High Court, District Court, Metropolitan Court. Any doubts? Hello? Okay. Now that is what is given here. It is the apex body of the judiciary, meaning the highest authority of the judiciary. It is established in 1950. Chief Justice is the highest authority. An individual can seek relief under Article 32 of Constitution of India. Meaning what, people? Under Article 32 it is given. If your fundamental rights are breached, you can directly come to Supreme Court. Where is it written? It is written in Article 32. Sir, can I go to High Court also? Yes, possible. Where is it written? It is written in Article 226. So remember, if your fundamental rights are breached, you can either go to Supreme Court or High Court. If you want to go to Supreme Court, it is written in 32. If you want to go to High Court, it is written in 226. Is this clear? High Court is the highest court of the state. High Court has three powers. One is called as appellant power, original power, supervisory jurisdiction. What do you mean by that? High Court has three powers. One is called as appellant power, original power, supervisory. What is this? Original means people. Under Article 226, people can directly come and file a case with me. Agreed? That is its original power. Directly it can take up cases. What is the second type of cases that a High Court can take? First, people will go to District Court. If they are not happy, they will come for an appeal. That case will come to me. That's the second power. That is only called as appellant power. That's originally someone directly coming to me. Appellant means people, something coming with appeal. Third one is called as supervisory. What is supervisory? There are so many districts in Karnataka. Agreed? In all the districts, there are courts. Who will regulate all these courts? There should be someone above all of them. Who will supervise? High Court will supervise. If you have filed a case in one district, but technically you should have filed it in other district, the Karnataka High Court will come and say, hey, why did you file it in that court? Da? You should technically go to this court. They will take the case from there. They will put it in the right court. That power is there with the High Courts. That's the third power called as supervisory. Is this clear, all of you? All of you? Yes. Chances of High Court is more. Remember and go. Clear, all of you? This is your judiciary. This is your first chapter. Any doubts? Hello? I hope it is clear. You tell me any doubt, I'll take up the doubt. If no doubt, we can go forward. Ministry of Law and Justice takes care of the implementing, and imagine tomorrow if there is any cases filed against the government, against the ministries, any of the government bodies. Now, how to regulate these entire cases? Who will fight? How do we have to take care? Who will pay? What will be the procedure? All that is given in that particular ministry. They will regulate. Public prosecutors. Now, for example, now I'll go and file a case. Now, for example, 2 months back, there was a case that was filed that one person fell because there was a pothole in the road. She was driving a bike. She fell and she has injured. Now, she wants to file a case on the government because of lack of roads. Now, who will come and fight? What is the entire procedure? So, it will all be governed and regulated by this particular ministry. Clear? Any other questions you guys have? No? Clear? All of you? 6 marks, pakka, remember and go, you will definitely get. And wherever I told you to remember, remember and go. You will have a question. Huh? Huh? Common law. Common law, any case can be an example. For example, Balfour versus Balfour can be an example. In the case of State of Delhi and Mukesh and others can be an example. Common law can be civil as well as criminal. Any case which is already decided and similar thing happens will be a common law. Yes. It can be civil as well as criminal. Any other questions? No? Done? Okay, that's your first chapter. Let's Indian Contract Act. Okay, this will take 1 hour. We will do one thing. We'll go for a break and come. Go for a break and come. Go. Have a good breakfast and come, and then we'll sit. Yes, So, what is the you're going for a breakfast break or how? Breakfast break? 30 minutes is good. Okay. Go for 30 minutes. Come back. Yes, people. Let's start with chapter 2, Indian Contract Act. Let's start the first unit. Nature of contract. Online audible done. Okay, back all of you. Okay, see here. Let's start with chapter 2, Indian Contract Act, Nature of Contract Act. Yes, we will. So, in Indian Contract Act, again, first chapter is nothing, it's just an introduction. Everything will come in Unit 2, Unit 3, Unit 4. But whatever is there in Unit 1, we'll see that. So, Unit 1 starts with what, people? Something called as essential conditions of a valid contract. What are the essential conditions of a valid contract? Yes. Concentrate. Dana, dosa, idli, kate, alla dana. Okay, now concentrate. Now, what are the essential elements of a valid contract, people? It is coming in two places. They have classified it into two things. One is something given under Section 10, something which is not given under Section 10, but which is still important. Yes? Okay. First, let us see something which is not given under Section 10. Now, what is that? The first one is, people, there has to be two parties involved. Now, it can be a natural person, it can be artificial person, but there can never be only one party. There should always be two parties. Next one is there has to be an intention to create legal obligation. What is this legal obligation or legal relationship? There is a case law here. What is the case law? Balfour versus Balfour. But what do you mean by intention to create legal relationship? In a simple word is nothing but at the time of entering into a contract, does the parties have an intention to take this contract commercially? What do you mean by that? If at all the other party does not perform the contract, I will take an action against him. I will take him to the court. Does the parties have that intention at the time of entering into a contract? For example, now you guys have paid some money to ArivuPro to join some particular course. Let us imagine money is taken, but the class is not made. We call up the class. Now, what is the first thing you guys will do? You guys will raise a ticket. You guys will raise a complaint. All that is done, but your issue is not solved. What do you guys do? You guys want to take revenge. Hey, how can these people do that? You guys do not mind going and filing a case in the court so that you can recover your money along with some justice. Now, while we are entering into these contracts, at the time of entering itself, we both are very clear. What? If I do not deliver, you are not going to compromise. If you do not pay, the academy does not compromise. Now, this intention is clear at the time of entering into the contract itself. Correct? Now, this only is called as what people intention to create legal relationship. What is legal? Legal is nothing but you have a right over the other party. If they do not do it, I will get it done. Now, let us imagine same thing. Let us imagine there is a person. Let us imagine. Okay, there is a housemaid who is working in our home. Now, you have promised your housemaid that I will take care of your children education. You have promised. Now, accordingly, the housemaid believed in you and the housemaid worked for you for the next 6 months thinking, yes, you will take care of the education. But you ended up saying that, so sorry, I cannot take care of your children education this year. Now, the question is, can your housemaid file a case on you for not living up to your promise? Because offer was there, acceptance was there. Now, can your housemaid file a case on you? No. Yes or no? Yes. How many of you think yes? Yes, exam question now. No? Someone is feeling yes and you're still feeling no, I should not raise my hand. Yeah? Now remember people, this is the difference. I told you, husband and wife, you always remember in law, you guys will understand examples. Yeah? This is exam question. Now, can the housemaid file a case on you? Answer is no. It's a domestic. Domestic is nothing but social agreement. Yes, it's an informal agreement, and it's not coming under charity. If you take charity also, then the question will come: what? Now let us imagine if charity has to come into picture in unit 2. I will give you a little more broader perspective about the same concept. Yeah, but these are called as what? Social agreements. Your friend telling you that I will file your IT returns, and your friend will not file it for you. Can you file a case? Answer is no, because you do not have that intention with your domestic people. Now, you and me, are we related? No. Now, when we enter into a contract, these are commercial. That's the difference between domestic contracts and commercial contracts. In commercial contracts, legal intention is proven. It is by default there. In domestic contracts, legal relationship won't be there. So, for example, a father promising their child that if you clear CA, I will give you a bike. The child worked really hard. The child cleared CA, but the father did not give a bike. Can the child file a case? See, because you guys are thinking from father and children perspective and you're saying no. Then what happened made in the CA case? That's what I say. You guys will just see the examples. Okay, father, okay, friend, okay. Maid comes, gone. Examples alone we will understand. Try to understand the intention. Are you getting the point? All of you? So in this case, what happened? The promise was serious only. But because they are a domestic contract, they are known people. They do not have the intention, oh, if my father does not give, I'll take him and file him in the court. You have all that intention? Say no at least, yeah. So we do not have that intention. But whereas in Arivu, you guys will say yes. If class is not done, you will go to court. Commercial intention is proven. That is what is called as intention to create legal obligation. Hello? So two known parties can never enter into a contract? Can they? How? Two known parties can never enter into a contract? They can? How? So now you will write in what is that? Consideration, exceptions, quid pro quo. There you will write what? Natural love and affection. It has to be registered. It should be in writing. Then you are proving hey, without intention, why will I write and get the instrument registered? I have intention now. That is why I'm going and getting the instrument registered. I'm paying some money. Now I'll rate, yes, there is an intention. So remember, that is the difference. If it's an unknown person, it's a commercial contract. Even without the instrument getting registered, there is a contract. It's a commercial contract. You have a right to file the case on other party. Whereas in a social or domestic, you will not by default get a right. You need to prove your right. How will you prove? Write down the instrument and get it registered. Exam question important. Clear on? Hello? Okay. Balfour versus Balfour is the case law here. Next one, other formalities to be complied. What is other formalities to be complied? For example, if there is, okay, there is a contract between you and me. You wanted to buy the class of Arivu and we were okay to give the classes to you. Now, this does not come under any other act. It is only governed by Indian Contract Act. So, we will follow only Indian Contract Act. Let us imagine there is a person who wants to buy a insurance policy. Now it's a contract again. I will give money, you will give me a policy. It's a contract again. I will follow Indian Contract Act. Along with Indian Contract Act, people, because it is insurance, insurance laws will also apply. Insurance Regulatory Development Authority, their laws will also apply. Now, according to them, if insurance contracts are to be valid, it should be in writing. But according to Indian Contract Act, a contract to be valid, it can be oral or in writing. No. So, if a contract is involving any other act, you have to satisfy the other acts as well. That's the meaning of the third point. Is this clear? Hello? Pakka? Okay. Next one, certain. What do you mean by certain? Tomorrow, your marathon starts. Which subject we will not tell. Okay, no, certain means what? Your contract has to be complete. It should not be vague. I want to buy 100 liters of oil. Which oil? It has to be certain. Tomorrow I will show you that movie. Which movie? It should be certain. So that is the meaning of not vague. If the contract is vague, then people, the contract is not valid. It is void. Is this clear, all of you? Okay. Next one, sir. Possible to perform. What do you mean possible to perform? It should not be impossible. So, for example, black magic. You come and do, let us do an Homa. We'll all pass CA. Yeah. So, all these are impossible to perform. So, on that, if you guys are believing in contracts, then the contract is void. Clear, all of you? So, these are certain things which is not there in section 10, but still they are important. Clear? Now, sir, in section 10, they are specifically given. There are certain things which is important. Section 10, that means it is given in the act only. Now, what is that? The first one is people, offer and acceptance. Second one, free consent. Capacity of parties, consideration, lawful object, not expressly declared void. Consideration, unit 2, we will see there. All other things, unit 3, we will see there. The first one is offer and acceptance, we'll see here. Clear, all of you? Okay. The first one, sir, is okay. Offer. Before that, okay. Before that, we'll do all these types of contracts only. Types of contracts, sir, depending upon the validity or enforceability. Very, very important. Again, students will go wrong here. Difference-based questions can be asked here. Remember, focus. The first one is called as people valid contract. Next one is called as people void contract. Next one is called as people Voidable contract. Next one is called as people. Illegal. Illegal contract can never exist. It can be illegal agreement. Yes, sir. Valid contract, voidable contract, illegal agreement, and void agreement. Unenforceable, we'll see. Now, what is the difference between these five? What is valid, what is void, voidable, illegal agreement, void agreement? Remember, Macha, if at all there are two parties, and if they have entered into offer plus acceptance, if they have satisfied the section 10 and not given in section 10, everything is satisfied. There's a tick mark here, there's a tick mark here. Then people, we call such things as a valid contract, and that is what is your definition. What is a contract definition? An agreement which is enforceable by law. What is agreement? Offer plus acceptance. When will it be enforceable by law? When you satisfy all the essential elements. So when an offer plus acceptance, that is when an agreement is enforceable by law, it is called as a valid contract. It's a proper contract. Done simplest form of contract. The next one is called as people void agreement. What is my void agreement? Sir, there is an offer. There is an acceptance. That means an agreement only. Sir, but it is not satisfying the essential elements of the contract. Example, sir, there is an offer, there is an acceptance, but it is with a minor. Is it a valid contract? Can you go to the court? Can you go to the court? Can I go? No. Then I have to give some name no for this. What is the name given? The name given is void agreement. Now you guys casually used no illegal contract. You can never use because once you call something as a contract, that means it is valid. Illegal means it is invalid. How can you club these two? Illegal contract can never exist at all. It is always to be termed as illegal agreement. The moment you call something as a contract, that means it is legal, it is valid. Only then it is called a contract. That's a logic. So void agreement means what? It's invalid, but still it's an agreement. But it is not protected under the law. Example is offer plus acceptance, but it's a minor. Agreed? All of you, it's called as a void agreement. Next one, let us take illegal agreement only. What is that? Sir, offer plus acceptance is there, but for what? Sir, the offer plus acceptance is given to go and kill a person, to drop a bomb. Sir, terrorist. Sir, we have given money to one person to go and drop a bomb in Delhi. Now, this is called as what? It's an agreement only. Of course, he has agreed with someone. But is it enforceable under the law? No. Now, this is called as what? Illegal. Why? Because it is not lawful. It is not lawful. Now, that is how it will become a illegal agreement. It's an agreement only, but it is punishable under the law. Hello? Yes? Okay. Next one, people. What do you mean by void contract? What is void contract? What is void? Void is void. Ceases to be enforceable by law. Like
certain things in the contract become mostly used
okay, right? Like as you guys said, right? Yes. So what is ceases to be enforceable by law? It's a valid contract. That's when the word contract has come. It is valid. So first it was very good. Everything was going good, but later it became invalid. Now, a contract which is initially valid, later on becomes valid. I mean, initially valid, later on it becomes invalid. It's called as people void contract. It is also called as supervening impossibility. Look at the names used. Supervening impossibility. Void contract. What are the reasons why a contract becomes void? Reasons. First one is supervening impossibility only. Next one, destruction of the subject matter. Next one is change of law. All these are the differences. These are the reasons why a contract will become void. Example of void contract, people. There was an offer, there was an acceptance, but there became a change in law. Sir, what do you mean by that? Sir, India-Pakistan match was going. All of a sudden, there was the attack between India and Pakistan. Immediately, India passed orders going forward until the government gives an order. Any contracts between Pakistan will come to an end. Sir, when will this such things happen? Yes, people, 2008. I don't know if you guys know. Shoaib Akhtar was playing for KKR. He's a Pakistani player. Shoaib Malik was playing for Mumbai Indians. Sania, what is it? Sania Mirza's ex-husband. He was playing for Mumbai Indians. Shoaib Akhtar was a fast bowler, Pakistani fast bowler. I hope you guys know. So he was playing for KKR, Kolkata Knight Riders, until 2008-9. Until then, there came a law which said that no, going forward, no, we cannot do anything with Pakistan. That is the day India has last played in Pakistan. Macham, recently Asian Cup, Pakistan hosted, but power of country. Just because India came to finals, the match only shifted to Dubai. Power of money. BCCI bigger than ICC. If you and why will ICC? Why do they have to listen? This will not be given to everyone. If other country is not interested, they will say, "Don't come. It's okay. Go." If your country does not want to play in Pakistan, go. If any other country had this condition, no, they will say, "Okay, go home. We don't want." But what is so special about BCCI? Nothing. If BCCI does not come, whoever is telecasting those channels, they will not get revenue. Because where is the maximum viewership? India. The telecast rights people will not buy it. Hotstar will not buy it. If India is not coming. Nice, no? So, now these are agreements. So, government will drop a bomb. They will say, Macha, today it is valid. Going forward, invalid. So, if they pass a law from that day, till today it was valid. Shoaib Akhtar and KKR was good. The day they dropped the bomb, Shoaib Akhtar had to cancel a contract. He doesn't have a choice. A contract when entered was good. After that, it became void. Such things are called as what? Void contract. This can happen due to change in law, destruction of subject matter, or it can be because of supervening impossibility. Supervening impossibility means what? When we didn't, meaning eventually it becomes impossible to perform. Destruction of subject matter means what? For example, for these two people, A gave his bike to B to use for some days and give it back. What type of contract is this? A gave his bike to B to use it for some time and give it back. Bailment, correct? Sir, while B was using the bike, what happened? Earthquake came, earth separated, bike went inside, earth came back. Now, where is the bike? Even B is also coming and searching, where is the bike? Correct, no? Now, people, what do I call these contracts? The destruction of subject matter. There is no bike any longer. Then what is the contract between A and B? So, void contract. Contract will come to an end. Who is liable or not? We'll see when we're doing bailment. For now, that is the example. This is clear, huh? Hello. Pakka, that's a void contract. I hope void contract is clear. Initially valid, later on becomes invalid. The last one is called as voidable contract. What is voidable contract? Voidable. Void means invalid. Able means you can do it. It is in your hands. Whose answer? A contract which can be voidable at the option of one party and not the option of the other. That means, yeah. So there is only one party who can decide whether this contract should be valid or invalid. If it is at the discretion of one person, then such contract will be called as what, people? Voidable. Example, people, is free consent. You guys have seen, no? What is that? Now, for example, anyone has bike here? Anyone who came in bike? Anyone who came in bike? Okay. What's your name? Jiva. I will say, Jiva, if you don't give me your bike, I will not allow you for tomorrow's class. Jiva will say, sir, no, sir, I'll give the bike. Alva, no. Say yes, da. See, he agreed. He agreed with his own free consent. No. 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 What is this called? Why not coercion? Jiva. No. What is this called?
You are in a position to Change dominant.
So
Dominant is feelings.
there is a relation. That is, he is a student. There is a teacher. Whenever there is a relation, coercion comes to an end. Undue influence opens up. And what did it? I said just Jiva. I didn't do anything else there.
No physical.
There is nothing which is punishable under the law. Meaning, imagine I'll say Jiva. Now, people, this is punishable under the law. I will threaten him, Macha, I'll kidnap you. Yes, sir. Jiva is like, yes, sir, you part-time gunda. Huh? Now, people, now this is what it's a threaten. Now it is punishable. There is coercion, undue influence. There is always a relationship, and one person should always be in a superior, dominant position. One person in an inferior position. Now, Jiva is in dominant, me in inferior. Student is always dominant. Hey, you also know that. Simply, Bernal. These are not simply. Society says teacher is superior. Where, da? In college and all, is teacher superior, ada? Hey, I know so many teachers da, who say, sir, bhaya sir, we feel scared to tell anything to students. Huh? And simply law says, oh, yes, teacher is superior. Where, da, macha? They'll take bubble gum and all and put on the bike seat itself. What and all they'll do, da? Huh? Huh? That and all they'll do. Now, people, now that is called as undue influence. Correct? No. Now, I took one blank document. I made Jiva sign. I took his bike. I will go to the class above and I took the bike from Jiva for 20,000. I'll go above for first floor. I will sell the same bike for 60,000. Everything, documents and all is in my name only. Now, do they know the story? You guys know because you have seen it. Do they know? No. For them, it's a valid contract. For you, it's a void agreement. So for them, it's valid. For you, it is void. So a contract which is balancing between void and invalid becomes what? Voidable. Now it all comes to what Jiva wants. What do you want, Jiva? My bike. Now Jiva says, sir, I want my bike back. Now if he comes and tell me, I'll definitely not give. He needs to go and tell it in a place where the difference happens. That is court. So if Jiva goes and registers a complaint, the court authorities will bring back, they will investigate the issue and they will take the document whichever he has signed, they will tear it. So a contract which looked valid on the face after tearing became invalid. That's why we give a name called as voidable. Jiva, it is your choice. If you want, not me, if you want, that is why it is called at the option of one party. It is his option, not mine. If he wants it, he can make it invalid. If he wants, he can make it valid also. What if he doesn't go to the court? It is a valid agreement. World will never know that all of this happened. Like the first floor. Agreed? That is only called as voidable. Important exam point of view. Remember and go. All five important. Clear? All of you? Okay, done. Next one. What is the unenforceable? Unenforceable. So a contract which is valid, but it has technical mistakes. Now, for example, correct? Jiva corrected? Correct. This is the example. Now, if I say Jiva, this is also Jiva only. But that Jiva says that is some Jiva, that is not my Jiva. It is not me, he says. Yes or no? Now, this is what is technical mistakes because in an agreement, name is important. If name is wrong, you can say, go and catch him, not me. So this is called as what? Unenforceable contracts. Clear? A contract is complete, but it has some technical mistakes in it. It's called as what? Unenforceable contracts. The next one, people, based on formation. This was based on validity or enforceability. Next one, based on formation. A contract can be further classified into. One is called express contract. What is express? Which is express. Dumbsharats banbadto. Huh? No, dumbsharats. Express means this. Implied means like this. You Express ನಿಮ್ನೆ ಕೇಳ್ಬೇಕು. What is express? Doubt ಆದ್ರೆ we'll see law now. Communicated verbally or written form. So whenever the terms and conditions are agreed, it can be oral or written. But how did you guys agree? I said whatever I want, whether in words or in writing, but I've communicated. You also have communicated what you want. When the parties have exchanged the words and then entered into a contract, it's called as express contract. What do you mean by implied? Implied, we are not speaking really here. Then we are just entering into a contract based upon conduct. The best example is your bus stop. The bus will come and stop, stand in front of you. You will just hop in. Gone are the days where they shout, majestic, majestic, Kormangla, Kormangla. Now they don't scream. You think you see the route, it goes to your route, you just hop in. Yes, when the bus stops near you, it's an implied offer that if you get in, I'll drop you in the desired place. The moment you step inside, it's a acceptance. It's an implied acceptance. Agreed? And remember always, there is something called as tacit contracts. What do you mean by tacit contracts? Silent contracts. There is nothing that you are speaking. Again, based upon conduct. The best example for tacit contracts is ATM machines, weighing machines, your vending machines. You drop your what is that? Coke can. That is also coming under this only. There is no one speaking there, but you are still entering into a contract. All of these are examples for tacit contracts, silent contracts. You're not speaking anything, but still there is a contract. What will you do? You put a coin, but that doesn't come. What do you do? First silent button I hit, sir. It will come. I know half the problems in India is fixed by hitting, but after that it doesn't come. Innೊಂದು ಕೊಡ್ತೀನಿ sir. At least somewhere you will call, Noda. Some after 15 times hitting, at least you call now. That is what they're telling you. You get a right. There is a contract. Agreed? Next one is called quasi. We will see when we are doing the unit only. Next one is called e-contract. What is e-contracts? The electronic contracts. Contracts entered over a digital platforms, electronic form. It's called as e-contracts. Example, Amazon, Flipkart, all those things. Next one is called as executed contracts based on performance. A contract can be classified into executed contract. Executed is nothing but past, done. A and B agreed. A agreed to deliver classes. B agreed to pay money. Classes delivered, money paid. That's all done. Next one is people executory contract. A agreed to deliver classes. B has paid money. You paid money on January 1st. But the classes happened till June. That is called as what? Executory contract. Executory can be two types. One is unilateral, bilateral. Unilateral is one party is pending. His job is pending. So, for example, in our case, if you paid the fees on day one, but we deliver the subjects for 6 months, so we come under unilateral executory contract. One party's performance is pending. What do you mean by bilateral? Both of us say, now I will say I will pay in, I will deliver in 6 months. You will also say, sir, I will pay in EMI. We both agreed today. Contract is entered today. But your obligation is also in future. My obligation is also in future. Then we call it as executory contract. Remember, in executory contract, we always exchange promises, not the product. In executed, product is exchanged. But in executory, promise is exchanged. I am promising to pay in future. I am promising to deliver in future. Understood? Yes, sir. So executory can be further classified into unilateral and bilateral. I hope this is clear. Any doubts? Hello? Okay. Next one, let us start with the essential elements of valid contract. The first essential element is offer. The first one they are telling you is classification of offer. Offer can be classified into express or implied, whatever we just saw. Next one is general offer. What do you mean by general offer? General offer is an offer made to public at large. So when we say big billion day sale, anyone can come and accept. CA registrations open from this day to this day. Any person eligible can register. So when an offer is made to public at large, anyone can come and buy. That is called as what people a general offer. Now in general offer, remember, there will be no express acceptance. You following the terms is called as acceptance. For example, you want to register for CA. You will not call ICA and say, sir, I have registered for CA. Are you happy? You will not say that, right? You will just file your marks cards, whatever is the required thing done. So you're just following the manual. Whatever they have said, you are following. That's all. That is only called as registration. There will be nothing that is acceptance in oral or in writing. Agreed? So remember always, in general offer, there will be no express acceptance. Case law here, Carlin versus Carbolic Smoke Oil Company. What happened? One company came and said, there is so much of COVID all around. If you use our tablets, you will not get COVID. Yeah. But one person took these tablets but still ended up getting COVID. Now this person wanted to file a case. Hey, COVID came down. What to do? That person said, see, there was an offer that if at all you use our tablets, that is medicine, you will not get COVID. But if you get, we will give you 500 rupees as reward. We have said, we gave an offer, but did you accept? Did you call it and say, I accept the challenge? Did you say that? Did you reply to our Instagram ad? Did you reply to our TV ad? No, no. Hello. When you have not accepted, then where is contract? Offer plus acceptance is important. No. Then so remember, here acceptance is not required. In a general offer, you take tablet, drink, that's all. That is only called as acceptance. You following the manual, prescription, whatever you are following, that itself is an acceptance. Here, so in general offer, there will be no acceptance. You following the terms itself is an acceptance. That is what happened here. And a person who was affected by influenza filed a case against the company, ended up getting the reward because general offer does not require any specific acceptance. Following the terms itself is an acceptance. Next one is specific offer. What is specific offer? Offer made to a specific person. A makes an offer to B, and who should accept it? B only should accept it, and that type of offer is called as people specific offer. If C accepts it, it is not a valid contract. Is this clear, all of you? Yes. We'll do one thing. I'll tell you here the case laws towards the end. I'll try to record all the case laws that is there in the book. I'll try to make that as a separate video. Yes. Try to watch it. It will be important. Yes. Okay. Only case laws. Let's try to cover that. Hello? Okay. So what is the case law for here? Specific offer. Moulton versus Jones. If you remember. Anyways, we'll take it up towards the last. Everything in one place. Okay. What is cross offer? Identical offers. Exchanging. A says that I have a car. Red car. I want to sell it for 5 lakh. Do you want to buy? Without being aware of this, B also writes one letter to A. I want to buy one car, your car, red car. The maximum I can pay is 5 lakh. Both of them exchange the similar offer. Now, is this a valid contract? Answer is no, because both of them have asked questions only. No one has given a reply. Cross offer is never a valid contract. It is exchange of identical offers. So when you say, I want to buy a car, and you say, I want to sell a car, without being aware of each other's offer, this will never result into a valid contract. So cross offer never leads to a valid contract. Next one is called as counter offer. What is counter offer? Exam important. They'll ask you counter offer scenario based questions. What is counter offer? Counter offer is also called as qualified acceptance. What do you mean by counter offer? For example, if our father goes and buys any vegetables, there is the vegetable Anna. Father asks, how much 1 kg of potato? Vegetable Anna says 40 rupees. Father gives 50 rupees. Ange will take potato, goes back. Valid contract. Now, mother goes, Vegetable anna, how much potato? 40 rupees. Mother, 4 rupees kurtiya. This is only called as what people? Counter offer. Counter offer is, hey, who cares what offer you give it? My offer is this. And the beauty of what mother does is what? You don't have an option also. It's not like a 4 or no. Hey, 4 only. You don't have an option. You have to give up. Yes or no? Now, people, this is only called as what? Counter offer. Now, salesperson is not giving the offer. Mother is giving the offer. Who should give acceptance? Sales guy have to give acceptance. Correct? No? This is only called as what people counter offer. Counter offer in a polished English language can also be called as negotiation. Wherever you negotiate is called as what people counter offer. If you guys watch Shark Tank, there you will see what is it? Counter offers. Yes, that's where you see counter offers. Okay, Bidri. Next one is called as standing or continuing offer. What is my standing or continuing offer? Offer which is standing is called as standing offer. Which is continuing is called continuing offer. What is continuing offer now? An offer which is open from certain time, 1st of Jan to 10th of Jan. Such type of offers is called, which is going on, continuing for a particular period. It's called as what? Continuing offer. People now think here, see here. There is a person called A. A gave an offer saying that I would want to sell my car and the offer is given today. You have 10 days to give me a reply. It is given on 1st of Jan. You can reply to me by 10th of Jan. Yeah. I followed British method. Okay, now. Okay. Now, people, you have 10 days time. I have clearly said in my offer, you have 10 days time. But people, by 5th day, I got a better offer from C. B has not yet accepted because he thought I still have time. But A people got a better offer from C and A accepted the offer. Now B is filing a case on A, saying it's a breach of contract. Now A has come to you and asking, dear students, is it a breach of contract? What is your answer? Is it a breach of contract? How many of you think it's a breach of contract? They lifted sir. Hey, yes or no? Lift. Is it a breach of contract? It's not a breach. How many of you think it's not a breach of contract? Hey, others so bought less. Not a breach of contract? It's not a breach? No? They think CA exam, ICA. They will tell your registration will be open from 1st to 10th. 5th only they will close the registration. Now, oh sir, your breach, injustice, sir. We'll go for strike only.
Can be revoked before the acceptance.
Offer can be revoked before the acceptance. Okay. See, remember, most of the people in exam, they wrote people, it's a standing or a continuing offer. And if A revokes it on the 5th day, it is a breach of contract. 70 to 75% people wrote that answer. The answer is no, people. It is not a breach of contract because acceptance is not done. And the last topic in first unit, what? Revocation of offer. If acceptance is not given, I have a right to take back my offer. Who cares whether I said 10, I'll give 15 days also. I will take back my offer. If you have not accepted, I think the terms have changed. I will take it back. That is okay. It is a revocation of offer. If it is not accepted, I can give a notice. I can revoke it as it is valid. Hence, it is not a breach of contract. Hello? Yes? Okay. Exam question. So, offer which is allowed to remain open for acceptance over a period of time. It can be taken back. Withdrawing is possible, provided it should not be accepted yet. Okay. Next one, communication. Okay, rules. What are the rules of valid offer? Maunam sammati lakshanam valid offer. Illa. Okay, valid offer. Okay. Essentials of a valid offer. First one, it must be capable of creating legal relationship. Balfour versus Balfour. Correct? Huh? It must be certain, definite, and not vague. 100 liters of oil. Which oil? It should be certain. It must be communicated to the offeree. Lalman Shukla versus Gauridhar. So A wants to sell something to B. This has to be communicated to B. If it is not communicated, of course, it is not a valid offer. Same way, if B says yes, it has to be communicated to A. If it is not communicated, even that is also not a valid acceptance. Both are important. And remember, offer has to be communicated same way. Acceptance also should be communicated by the person who has the right to communicate. Someone cannot communicate. You guys should have seen your exam-based questions. That school, a teacher would have applied for a job in a school. The teacher has a friend in the school who said that your role is almost selected, but she gets a rejection offer. Now the teacher wants to file a case on the school saying that I knew that my candidature was selected, but I got a rejection email. So it's a breach of contract. The teacher wants to file a case. The first thing here, the friend gave you a hint that your candidature is selected. Is it a valid acceptance? No. Answer is no. You have to get acceptance from a formal, official person who has a right to do it, not from a random person. Correct? Huh? Yes, sir. That question you guys would have seen. Okay, next one. It must be made with a view. Again, case laws will do at the end. It must be made with a view to obtaining the assent of the other party. Meaning, you have to give the other person a choice to say yes or a no. If you say it as a command, it can never be an offer. Yes, sir. Now, Shivgami told Katappa to go and kill Bahubali. Did he have a choice? It's not an offer. It's an order. Correct? Now, it may be conditional. You will get a free delivery. Flipkart provided your cart value is 500. Offer can be conditional. So first, if you want to get a free delivery, you have to first meet the condition of cart value. So offer can be conditional. It is valid. Next one, offer should not contain a term that non-compliance of which would amount to acceptance. Same thing. In short, people what? For example, I will write a letter. A writes a letter to B saying that I want to sell my car to you for 5 lakh rupees. You have 1 week to reply. If you do not reply within 1 week, that means I assume that it is an acceptance. Such things is not considered as a valid offer. So if B does not reply in 1 week, it will not become a valid contract. You have to give a choice to the other party to choose. If you do not reply, if you do not do that, it is an acceptance, can never be considered as a valid contract, is what they are telling you. Clear? Huh? Okay, next one. Offer is different from mere statement of intention, invitation to offer, communication. What is the offer is different from invitation to an offer. Important, very, very important. Offer is different from invitation to offer. What do you mean by that? What is invitation to an offer? Inviting a what is invitation to an offer? So, for example, people, you guys get a newspaper ad, you guys get an Instagram ad saying that if you guys come to the store on so and so day, then you will get all the products at 50% discount. Now, this is an ad, it's not an offer. If you guys are looking at it and if you're going to the store, now you actually go, you pick up the goods you want, you go and stand in the counter to bill it. Now you are making an offer. Now the cashier will take it. He will say, yes, it is eligible. It will come under the offer or not. He will tell. If it is not covered under the offer, then you will not get the offer. So in an invitation to offer, always remember the salesperson will give you an invitation. Why is this invitation for? He's giving you an invitation to please come and make an offer. You make an offer. So always remember the buyer makes the offer. Then what does the salesperson do? The salesperson does a acceptance. Is this clear? Huh? Hello? Something. Yado not madi. Now see here. See this question, exam question. Ashok goes to the supermarket to buy an air conditioner. He selects a branded air conditioner having a price tag of 14,000 after discount of 30,000. 3,000, sorry. Ashok reaches at cash counter to make the payment. But the cashier says, sorry, sir, the discount was up to yesterday. There is no discount today. Hence, you have to pay 43,000. Ashok got angry and insisted for 40,000. State with reasons whether under Indian Contract Act, can Ashok enforce the cashier to sell at a discounted price? That is 40,000. Can he do? Understood all of you? So, add was, sir, please come in. There is a 3%, 3,000 discount. Invitation, you came inside. When you saw it, you took it. Of course, you do not know the terms yet. He said the discount has ended yesterday. So you took the air conditioner you want. You're standing in the queue now, the billing. You said, I want it for 40,000 as per the price. He said, sir, I'm so sorry. At this price, we will not be able to give. You are making the offer. I want to buy at this price. Can you sell? Now the salesperson has to say yes. If he had said yes, offer plus acceptance, contract is made. So here, what will I write? Remember, invitation to an offer is different from offer. Here, the salesperson giving an ad that there is a discounted sale is an invitation to an offer. The buyer willing to buy the product for 40,000 was an offer, where the salesperson has a choice to say yes or a no. Now here it was a no because the offer has ended, and hence do you have a right? Can Ashok, how will my answer be? First will be my provision. I will split my question, my answer into 3 paragraphs. My first paragraph will be the provision. What does the law say? Law, here do not put your brain. You have to put what is there in the book. Cut, copy, paste. That has to be your first paragraph. My first paragraph has to be here. Offer is different from invitation to an offer. In an invitation to an offer, the salesperson invites the buyer to make an offer and the salesperson gives an acceptance. So mere invitation to an offer does not have any binding effect on the contract. In the given example, whatever the salesperson did, it's a invitation to an offer. That's my provision. Now, second paragraph, in the given case, who is it? Air conditioner shop. Okay. Ashok goes to a shop. He selects a air conditioner and he is requesting for the price of 40,000. Now, that's a fact. Facts is given in the question only. Rewrite it. Remember, the lesser the facts, the better for you. Because you know, I know, the examiner knows. You're copying. Facts is nothing but whatever are there in the question. Take 3 points and write down as it is. So first paragraph will be my provision. That is clear. Second paragraph will be facts. In that I will write Ashok wants to buy the air conditioner 40,000 after a discount of 3,000. Second fact, the sales guy has informed Ashok that the discounted sale has ended yesterday. The matter of question is, can Ashok get the air conditioner for 40,000? Question mark. Done. My 3 facts. Now comes conclusion. Conclusion, don't use your brain at all. They would have already given it in the question. What is the last line saying? Can Ashok enforce? Answer is, can Ashok enforce? No. Rewrite the same thing. Ashok cannot enforce. That's your conclusion. And remember, conclusion should always be customized. Use the names. Don't use the names in provision. Use the names in the conclusion. So in my conclusion, I'll be writing that as the air conditioner guy has made an invitation to an offer, the air conditioner guy is not supposed to, or not bounded to sell the air conditioner at 43,000. Hence, Ashok cannot enforce the cashier to sell at a discounted price, as it was a mere invitation to an offer and not offer. You write a mancha, exam value will come and argue. Clear? Hello? That's how you're supposed to write exam question. Is clear? I hope something is going inside. So what I've done is I've taken some such little tricky questions and let us discuss that simultaneously as and when the unit is going. Clear? At least something will let us make some difference. Okay, that was the essential conditions of. Okay, anything else was there? Did I cover everything? Invitation to make an offer. Okay, and what is that? Statement of a price or intention or answer to a question cannot be considered as offer or an acceptance. Sir. We saw it in the case of what? Harvey versus Facey. What is that? In this case, what happened? A made an offer to B. I want to buy your bumper hall pen. Imagine land. A wants to buy B's land. So I wrote a letter. In that letter, I have 2 questions. What are the 2 questions? First one, are you willing to sell the land? Are you willing to sell the land? Second one is, what is the best lowest price possible? What is the best low price possible? Now the other party replied, B replied, the best lowest possible price is 1 lakh rupees. A said, I'm okay with this particular price. Now B rejected selling the land. A filed a case. Sir, I asked him a question. He replied, I said yes. Now he is saying I will not sell the land. Hence it's a breach of contract. The question is, in the breach of contract? No, because of 2 grounds. What is that? First one, just replying price does not mean that I'm interested to sell. Because the first question was clear. Are you willing to sell? He has not answered that. So remember, a reply to a question and just quotation, quoting a price cannot be taken as an offer or an acceptance. That is what is the case law Harvey versus Spacey. Offer is different, quotation of price is different, answer to a question is different. You cannot take it as an offer. Correct? Yes, sir. Hello, all of you. Okay. Next one is people, acceptance. What is acceptance? Rules of acceptance. William Anson's metaphor, will come back to that. Acceptance can be given only by the person to whom the offer is made. What is such acceptance called as? Specific offer, specific acceptance. It can be only, acceptance can be given by the person to whom the offer is made. Next one, acceptance must be absolute and unqualified. This is only nothing but qualified acceptance or counter offer. You should never be a counter offer. We should, meaning if mother goes, not valid contract. Father goes, valid contract. Remember that. Hey, don't judge me. Simply said down. Okay. Now people, correct? So wherever there is no negotiation, it's a valid contract. If there is a negotiation, it's not a valid contract. Agreed? Meaning when I say it's not a valid contract, offer will no longer be by the person whom it is made. So in our case, Tomato Anna made an offer that the tomato is for 40 rupees. But the counter offer is made by the mother. It is for 4 rupees. Now this becomes the offer. Then Tomato Anna's offer came to an end. Correct? Huh? Yes or no? So always remember, in counter offer always rejects the initial offer. When a 4 rupee offer is made, 40 rupee offer comes to an end. Agreed? Huh? Yes, sir. Okay. Acceptance must be communicated. Huh? Cross offer and counter offer both are not valid, you're saying. Counter offer does not form a contract at all. In counter offer, the first offer comes to an end. It will be replaced with the second offer. If you give an acceptance to that, that can be a valid contract. But in cross and counter, both in itself will not form a contract. Correct? Huh? Okay, the acceptance must be communicated. I told you offer also should be communicated. Acceptance also should be communicated. Brockton versus Metropolitan Railway Company. In case of, we'll look at the end. Next one, acceptance must be in the prescribed mode. What do you mean by that? If I've clearly told you, give me a reply in an email, you have to reply to me in an email only. So that is the meaning of acceptance in the prescribed mode. But remember, I have told you to give me the acceptance in the email, but you gave me in a WhatsApp message. Is it a valid acceptance? Is it a valid acceptance? Remember, the seller has to say that to the buyer, because it is not in the prescribed mode, I will not accept this offer. If it is not communicated, it becomes a valid acceptance. How many of you understood? How many of you didn't understand? They may ask you the exam. They may ask you a question in the exam on this point. A told B, if you are okay with the offer, give me your acceptance by an email. A told B, if you're okay with the offer, give me the acceptance by an email. But what did B do? B sent a WhatsApp message. Now, is it a valid acceptance? No. Now, what should A do? A should communicate the same thing to B. As I had clearly mentioned that the acceptance should be in email, you have given in WhatsApp, I will not entertain this acceptance. It's not valid because it is not in the prescribed mode. A has to communicate. What if A does not communicate? It will become a valid acceptance. High chance of question being asked. If it is not communicated, it becomes an acceptance, even though it is not in the prescribed mode. Understood? Hello? Now see, read it here. Read this point. Where the mode of acceptance is prescribed in the proposal, email. It must be accepted in the email. But if the proposer does not insist on the proposal being accepted in that manner, after it has been accepted in another manner, WhatsApp, the proposer is presumed to have consented to the acceptance and it becomes a valid contract. It is your duty to communicate. I'm not okay with WhatsApp. If you do not communicate, it will become a valid contract. On this point, they can ask your questions. Remember and go. Clear? Hello? Next one, time. Acceptance always has to be given within the given time. Next one is mere silence is not an acceptance. Maunam sammati lakshanam does not work. There has to be a specific, express acceptance or implied acceptance. But silence cannot be taken as an acceptance. What do you mean by that? A tells B, if you do not reply, I will assume it's an yes. Cannot be a valid contract. Yes? Okay. Acceptance by conduct or implied, anything is okay. It can be express also, implied also. You getting into a bus is an implied acceptance. Try to tell. They're asking you, whether the following does it constitute a valid contract? Take a guess. I mean, try to answer. J takes a seat in the public bus. Is it a valid contract? Yes, because it's an implied acceptance. J tells M that N has expressed his willingness to marry her. J tells M that N has expressed, you're not able to see. Only you're able to see it. Audible? Don't tell me. Okay, no. J tells M that N has expressed his willingness to marry her. Is it a valid contract? Why? Uh-huh. Acceptance must be communicated. Is it a valid contract? Marriage is a contract. Huh? Yes, sir. Marriage is a contract. Huh? Is marriage a contract? Is it? A tells B, I will marry you. B says yes. And A does not marry B. Can B file a case on A? Can B file case on A? This and all we can file a case. That is divorce. I'm saying here marriage did not happen. That is marriage done. This is marriage not yet done. Can A file a, I mean, can B file a case on A? Huh? It's a social contract. Agreed, huh? B can file a case on A. Macha, vindictive or exemplary damage. Vindictive or exemplary damage can be claimed only in two cases. One is wrongful dishonor of checker. Second one, failure to marry. Only in those two cases, vindictive or exemplary can come. It is there in a syllabus, not out of the syllabus. So, according to that, yes, it's a valid contract. Allah, but this all I'm telling my example. See, no. You've come. I will answer. Wait. Okay, see, one thing, whenever we are taking the facts, we are assuming that you can prove it. If I am not questioning or I'm not coming on the point, whether it can be proved, answer is yes, we assume. Imagine it can be an engagement, it can be a message, it can be a call, it can be a witness. So for example, in boys gang, one person is in relationship, the entire class will know. Witness, take everyone to the court. Yes. So how is always a matter of fact. But my question is, even if I prove, is it a contract? Answer is yes. Yeah. And I'm not saying out of the syllabus, that it is there in the syllabus. Exemplary. Macha, you know what is my vindictive word, you know? You guys remember reading the word vindictive damage, huh? The word vindictive means revenge. I want revenge. B, sir. So, you want to take revenge emotionally that this person has been invested in you. You can seek damage. And the word you need to write in your court's plaint is called as, sir, mental trauma. Yes, sir. Mental trauma. Yes, sir. See, in the instant case, there is no contract as an essential element of communication offered by one party and its acceptance by the other party is missing. Only one way it's there. Agreed? See, they are not telling a social, the domestic, that's why it's not a contract. Did they say that? No, it's a contract. Yes? How long? Who said? Tell me. How is marriage a contract is you saying? Here it is not a contract. Where did I say this is a contract? I'm telling you, A proposed B that will you marry me? B said yes.
It's a contract.
That only I said it. This side didn't tell it. Yarda me. That did I'm telling you. This is not a contract. That is a contract. Here there is no contract because there is no acceptance. Okay, na G. You're convinced.
Yes.
Okay. J bids at public auction. Is it a contract?
Sir.
Huh? J bids, bidding. Is it a contract? They said Tala 7 for a reason is for sale. He said, "Yanakku veno." Is it a contract or not? Yes or no? Just the bidding will not give you any right, people. You should win the bid. It should be a highest bid. All that will come into picture. Just giving your bid will not make you win the auction. You have to be amongst the competitive bid. Only then you'll win the auction. So it is not a valid contract until that's the highest bid. J puts three 1 rupee coins in the slot of a platform ticket vending machine at the railway station. Is it a valid contract? Is this a valid contract? Is this a contract? Yes, it is a valid contract. Tacit contract. Implied contract. Implied. A engages B to do certain that engagement Allah. A engages B. She's already speaking, sir. You leave this wedding to engagement and all. A engages B to do certain work and remuneration to be fixed by C. I say, you come and work. I will pay whatever he tells me to pay. A called a carpenter. I asked him to make a sofa. How much should I pay? I will pay whatever C tells me to pay. I will pay that much. Is this a valid contract?
Yes, sir.
Is it a valid contract? How can this be a valid contract? Huh? Is it a valid contract? Is it vague? It's a vague contract. It's a valid contract. Sir, how can you say, sir? It's a valid contract. I'll give you one example. Forget about Indian Contract Act. In Sales of Goods Act, a price can be determined by the parties themselves or by the valuer. You either seen it, Unit 1, ascertainment of price. Sir, the Sale of Goods Act. This is the Indian Contract Act. Say, in the class, I would have told you, Sale of Goods Act was first a part of Indian Contract Act only. So it's a continuation of the act. Yes, it is there in a different act today. But when Indian Contract was made, Sale of Goods Act was also part of Indian Contract Act only. So the price can be agreed by the third party, but both of us should be okay with it. Understood? But when we are doing that part, I tell you, A and B promise to pay for the studies of their mate's son. Valid contract. Social or domestic intention to create legal relationship is not there. A chartered accountant promises to help his friend to file his IT return. Commercial Allah. Correct? It's not a valid contract because social or domestic. Is this clear, all of you? Okay. Next, communication of offer and acceptance. When does an offer and acceptance come to an end? This is the rule. Hello. When is an offer complete? When is an acceptance complete? Offer is complete when offer is complete. Acceptance complete. When is offer complete? Lip sync fellows. How many of you know this concept? How many of you don't know this concept? Confused. Confused. Okay. People offer acceptance. When is an offer complete? When is an acceptance complete? A and B. A is there, B is there. Agreed? First assumption. Remember, if you guys have to understand Indian Contract Act really good, do not read it with today's technology. You guys have to believe this. You are in 1872. And the mode of communication is letters. Because remember, when this law was made, 1872, WhatsApp was not there. So the contract was written in a way that keeping letters in mind. So today you guys will think, well, sir, all this, how can it happen? Means, then what do I say? I have to convince you with an 1872 Act in 2025. So you have to read it as if you are in 1872. That doesn't really make sense. Clear? Okay. When does an offer complete? Meaning, when does offer come into existence? When is it considered as, okay, now offer is made to the other party? How? When is it complete? Communication of offer is complete when it comes to the knowledge of the person to whom it is made. A made an offer to B. Much I want to sell my car. Now B, when will it come to his knowledge that A has made an offer to me? Let us imagine I wrote a letter. A got the letter. A opened it. A read it. B reads it. Whenever B reads it is when he's getting to know, okay, it's an offer. B is not chitty robot. I got a letter, unge scan, I'll get to know what is inside and all. I have to open and read it. That's when I'll get to know. Now, people, that is what they're telling you. Whenever B reads it is when the offer is coming to an end. It is completed. Offer is completed. Now, when is acceptance completed? They're telling you. B wrote an yes. He posted in a post dabba. Yes, sir. Now, when is the acceptance completed? They're telling you, Macha, acceptance, when it is completed, it depends from two perspectives. From B's perspective, one. From A's perspective, two. So acceptance is complete. First, from B's perspective, when is acceptance complete? From A's perspective, when is acceptance complete? They're telling you. First, as against the proposer. Who is proposer? A. For A, when is the acceptance complete? They're telling you when it is put in the course of transmission. What do you mean by that? B took a letter. He saw A wanted to sell his car for 5 lakh rupees. B turned the page. He wrote, yes, I am interested. I've written my yes. I've taken, I've posted it, I've put a stamp, I've put it in post dabba. Now, can I take it back? No, don't tell us, sir. I'll put my hand, I'll take it. Legally, can you take it? No. Now, people, you have put the letter in the transmission, meaning the transmission, the process of transfer has started. The day you put it into that people, now A can no longer take back his letter. You remember, go back to the standing offer I told you. I told you that the offer will be open from 1st to 10th. Yeah. On 5th, B replied saying that I want your car. I have put it in my post dabba. Now A wants to take back his offer because A got a better offer for the car. Now imagine A wrote a letter to B. I want to sell my car for 5 lakh. Now on 5th, B accepted. He has put the letter in the dabba also, but A has not yet received the letter. But B has just put it in the post dabba. Now, people, on 6th, Mr. C comes and tells A, hey, can you sell me your car? It's a beautiful car. I'll give you 7 lakh rupees. Now, A wants to buy it because he's getting it at a better price. Now, you tell me, can A sell his car to C? Can he take back the offer made to B? No. The answer is, people, acceptance is complete. Offer was there. Acceptance is also complete. Even though A has not read it, B has replied to it. Done. A cannot take back the offer. It is done. Revocation is not possible. Why? Because against A, when is the acceptance complete? Whenever B puts the letter into the transmission, into the dabba, it need not reach. The moment I reply, that's the end. I cannot take back the offer because acceptance is complete. Is this clear? Hello? Next, as against the acceptor. Who is the acceptor? B. For him, when is the acceptance complete? When it comes to the knowledge of the proposer. Who is proposer? A. When will it come to the knowledge of the proposer? The letter has to reach A. A has to take it. A has to read it. Whenever A reads it, is when the offer acceptance is completed from the B's perspective. Hello? What do I mean by that? Now, when did B reply, people? 6th January 2026, B replied. Agreed? Now, sir, let us imagine on 8th Jan. Okay, let us imagine on 9th January, the post reaches A on 9th Jan. But on 8th Jan, people, Mr. D came and made another offer to B. Hey, why do you want to buy his car for 5 lakhs? The same car even I have. I'll give it to you for 3 lakhs only. I'll give it to you 3 lakhs only. Now the question is, can B cancel his acceptance? Yes. He has replied on 6th only. It will reach him on 9th. On 8th, can I cancel my acceptance? Can A cancel it? Can B cancel it? 100% all of you? Pakka? Remember, A cannot cancel, B can cancel because the acceptance has not yet reached A. It is not yet complete. From B's perspective, B still has time to take back his acceptance. How? I will write one speed post with a hope that speed post will reach first. Now let us imagine, on 8th I wrote a speed post. I do not want your offer. Now speed post also reached. That is, no also reached. Yes also reached. Which one will prevail? It depends, people. A, whatever he reads first will prevail. Now it's an assumption. I might read A. I might read yes, but I might say I have read no. It's an assumption that, okay, I'm reading yes only and I'm telling yes only. Is this clear? Exam point of view, they can ask you a question. Remember and go, important. Same thing, everything I've put here in the form of example. Take a minute, see it, if you guys understand. Kamakshi has a question. Why is it called as an Indian Contract Act when we got independence only in 1947? Aha. Huh? Hey, we got independence in 1947. Before that, you were not India, huh? You were India only. Hey, Bharat was in that history when king was there, huh? It is called as India for a very long time. Hey, in 14th century only were called as India. They did not call it as Independent Indian Contract Act. They called Indian Contract Act. And just for your information, Indian Contract Act does not belong to India because we did not make it. Indian Contract Act was made by Britishers. And just for your information, in 1947, we made one book. That book is called Constitution of India. We made in 1947. Implemented in 1950, that happened. Okay. Constitution of India has been amended 110 times. More than 100 times. Indian Constitution is amended. Indian Contract Act, which is written in 1872, is not even amended 3 times. An act which is close to 150-year-old is not even amended 3 times. That's the power of writing. Absolutely zero confusion. In the law, you know one thing, whatever examples you'll be seeing, those examples are not created by anyone. Those examples are written in the law by the lawmaker itself. No other law will have it. See, that's the beauty, no? Wherever we have to appreciate, we have to appreciate. Huh? Because we first say this is how it is. Later, it will not be logical. For example, Jammu and Kashmir, when it was written, Jammu and Kashmir did not belong to neither us nor to Pakistan. But with time, it changed. Now, if you see, old syllabus people studied Indian Contract Act applies to entire India except Jammu and Kashmir. But you guys are studying it applies to Jammu and Kashmir also. Because that time that was a law. Now it is different. Correct, no? That's what I'm telling you. Hey, India means it was India only, no, before also. You India. Okay. Understood? Hello, looks clear? Okay, the last ones are modes of revocation. How can I revoke my offer? First one is by notice. Macha, offer comes to an end. Done. Intimate and revoke it. Second one is by lapse of time. 10 days given. 10 days you don't reply. The offer comes to an end. By non-fulfillment of condition precedent. If you guys want Flipkart, free delivery, that means your cart value should be 500. If 500 is not satisfied, offer comes to an end. Next one, by death or insanity. I make an offer, but the person died. Of course, offer comes to an end. But we'll be seeing the extended version of it in the third unit. That time we will see. Next one, by counter offer. I told you, tomato anna 40, mother 4 rupees. The 40 rupees comes to an end. Correct now? Next one, non-acceptance in prescribed mode. Email or WhatsApp provided. Communication is very important. You have to say that it is not in the prescribed mode. If not, it will be a valid acceptance. Next one, subsequent illegality. What is this, sir? Initially, macha nothing but void contract. When you guys made, it was valid. Later on, Shoaib Akhtar, Pakistan became invalid. Subsequent illegality. TikTok, இருக்கா இப்போ இருக்கா இல்ல PUBG இருக்கா இல்ல why change in law subsequent illegality cam scanner app you know cam scanner is there no it's not there PUBG we play sir we are very clever anyone tell me your name I'll tell that this person plays tell me your name who plays PUBG hey, you'll play a PUBG tell me name see now got to know what is legal illegal tell me your name and you say that you will play PUBG agreed yes it is illegal you guys are doing it but it's illegal it's just like your share auto on a bike it is not allowed but you are doing it that's all so that's where subsequent illegality comes into picture is this clear all of you okay done any doubts that's your unit 1 okay next one unit 2 takadak legal rules regarding consideration what is consideration something in written is called as consideration quid pro quo quid pro quo okay legal rules regarding consideration it must move at the desire of the promisor what do you mean by that people if someone doesn't voluntarily it will never be called as a contract it must be move it must move at the desire of the promisor means I should have asked for it if you do it voluntarily it is never a contract any example for that it must move at the desire of the promisor ಮೆಡಿಟೇಷನ್ ಆದ್ರೆ ಆನ್ಸರ್ ಮೆಡಿಟೇಷನ್ ಮಾಡ್ಕೋಬಿಟ್ರು ಡೇ ತಿಳಿದ how to make the class silent by asking questions okay it must move the desire of the promisor day mancha you find one wallet last bench if you find a wallet what do you do depends I'll see first yeah no one then me only ಹಂಗೆ ಹಾಕೊಂಡು ಹಂಗೆ ಜುಟ್ಟು ಕರೆಕ್ಟ್ ನೋಡ no what do you do if you find a wallet Check? That's what. Check the money is there or not. Correct. He's a very sincere student. Yeah? Correct, Noda? Of course, all of you will do that only, no? See, boys accept it. You ask girls what they will say. Ask check. What girls, what will you do? Da? Sir, we will not take it. We will honestly go and give it to the owner. Or, sir, we will give it to the police station. Ask. Hey, what do you do, Tilda?
They could be common people do the same thing.
But what? But what did you say? Same as what? Sir, I will give it to the owner. Huh? Correct, Oda? What will you guys do? Da? What will you do? Da? Take little, sir. Full papa venda. Half papa. Huh? Karma comes back, sir. So let half of it come back. Not full. This ideological. Okay. Huh? Sir, no one should know that I took it. It should be natural. So, this is what people. Now imagine A got the purse. A went to B and said, yes, let us take your answer only. Girl's answer. Sir, we will search the owner. Now they searched the owner. They went and they gave back the purse also. And that person went. He took the purse. I mean, B, okay, let us imagine. A came to B's door. A said, sir, I found your purse. Please take it. B was like, oh, very nice. Thank you. He took the purse. He closed the door. So the girls are standing. Sir, cab. I came in cab. At least 500 rupees. You have to give me for the cab price, no? At least he has to take care of that, Noda. Cab or at least auto. At least bus. You have to give it or not. Now, people, the girl who came and returned the wallet is expecting for some money in return. Will she get it or not? Why? So the extended rights we will see, but this is only called as what people. We have not seen the complete one here. Quasi contracts will come. But people, it must move on the desire of the promiser people. That is the meaning. Did I ask you to come and give it to me? I will say, hey, I wanted to throw it there. Da. It was waste. I had extra. I put it there. Why did you bring it to me? Now, people, if I do it, if I'm doing it voluntarily, remember, people, I cannot get any right over it. But the extended version, I will tell you. Yeah. But for now, that is the meaning of this. When you do something voluntarily, you cannot expect anything out of it. Are you getting the point? Yes? Okay. Screen is not clear, voice is not clear. My half-life based. Nothing is clear. Now it's okay, yeah? Okay. It must move from promisee or any other person. What do you mean by that? Promisee or any other person? A, B, they are telling you whatever is the consideration, it can be given by A only, B only, or C can come and tell on behalf of A, I am giving. This is also considered as a valid consideration. I can only give it, or someone else can also give it on behalf of me. Chennai versus Ramu. What happened? There is no girl here. How? What is that? Correct. Chennai versus Ramaya case. What happened there? There is. Girl is not here. Ramaya. Okay, now you are convinced, huh? Happy, yeah? Sita, for your satisfaction, will change name also. What is there? You want girl there. Girl is there. Girl irka. எல்லாம் இருக்கு. Okay, now see here. Everybody see da. Now see da here. What is the case law of Chennai versus Ramaiah? Garla. What is the case law da? அவங்க preparation for exam இப்படிதான் இருக்கு. Brother and daughter, mother and daughter, they enter into a contract. Okay, there will be a old lady da. She will have land. Now I will tell. Now old lady will have a land. The daughter will ask, hey, what is it, mother? Can you please give me that land? The old lady will say, I give you the land, provided I have one of my brother who is equally aged as mine. If you take care of him every month, I will give you the land now. She said yes. She even said yes to the uncle also. She said, yes, I will take care of you. An acknowledgement was given. After acknowledgement, the mother transferred the land and she died. The lady became KD. She said, I will not give the money anymore. Now the uncle went and filed a case on this lady asking for the money. Now she said, there is no quid pro quo, hence it is not a valid contract. I am giving you something. What are you giving me in return? Now this uncle quoted something called AUKD. Remember, the consideration can move from the promisor or any other person. So whatever my sister gave, that is a consideration for my contract. Hence it's a valid contract. Consideration may be past, present, or future. We have already seen this in executed and executory contract. It need not be adequate. Remember, they'll ask a question here. What do you mean by need not be adequate? This pen costs 10,000 rupees. I want to sell it away for 100 rupees. Anyone wants? Anyone wants? Anyone tell da? Anyone wants? Ase. Ase. Anyone wants? Okay. Now, people, this is only called as what? Consideration need not be adequate. The value is 10,000. I need not sell it at the same price. But this will not affect the validity of contract. Tomorrow I cannot only come and say, hey, how can I sell it for 100? 10,000 worth product. So you cannot question the validity of the contract based on price. Even if it is 1 rupee, it's a valid contract. If it is 0, is it a valid contract? I'll give this product for free of cost. Is it a valid contract? Is it a valid contract? No. Why? Quid pro quo is a valid essential element. So free, no. 1 rupee, yes. Diagonally also. Okay. Performance of what one is legally bound to? Understood? What is this? Performance of what one is legally bound to perform. Now, for example, what is your name? Nitish. Nitish is going on road now. One police uncle will stop your bike. What will the police uncle do? Tell me. He'll ask for driving license. Do you have a LLR? Okay. Were you wearing helmet or no? Say no. No. Now he catches you. What will he do? Tell me. Fine only, no? Tell la. Huh? Yeah, no, Indian also. What? Tell la only da. What is your name? Sir, no, sir. Name and friend, sir. Hey, bribe is there in our system. In India, bribe is there. Bribe. Where? Where? Tell me 1%. Name, I'll take name and I'll write bribe. Silent. Okay, according to me, I don't know. There is no bribe. Anyone thinks there is bribe? Tell me. What is your name? Tell me. Alba. So you also tell the same thing. There is no bribe. Like we have said it to all other Indians. Correct? No? Okay, now see here. Performance of what one is legally bound to perform is that, people. What is that? It's your responsibility. Let us imagine Okay, now listen. If a cop is solving a case, but the cop is expecting something in return, can he expect? Answer is no. That is only called as performance of what one is legally to perform. You cannot claim it as a consideration. For example, doctor says, now, for example, imagine, sir, you have a complicated open heart surgery to be done. We have to remove the kidney pipes and all. We have to do welding. It takes time. So we charge 5 lakh rupees for this operation. After operation, the welding was successful. The patient is alive. Now people, the doctor charges, sir, you're alive, so we will charge 5 lakh extra. Can I charge? Why? You're not happy that this person is alive after welding? Then that is only called as performance of what one is legally bound to perform. That is your duty. You cannot charge extra again. Lawyer cannot say, I will fight your case. If I win, I'll again need extra money. You will get your money for fighting the case. That is for winning only. You cannot say, if I win, I'll get extra money. One example question, that firefighter. One day, what happened? One place full of fire. Full. Yes, sir. Full fire was there in one property. So one uncle called a firefighter. Fire engine, da. So the fire engine, one lady came. One lady came and she put off the fire. She put off the fire. Now this uncle came and said, okay, this lady went and asked, sir, how was this? I did it. Okay. He said, okay. Sir, can you give me 10,000 rupees? Uncle said, okay, come tomorrow. Tomorrow this lady went, but this uncle did not give this 10,000 rupees. Now this lady wants to file a case on him for recovering this money, which she gave an offer 10K. He said, okay. Now people, she's not getting that 10K. So can she go and file a case on him in the court? Yes or no? Offer was there, acceptance was there. Can she file a case on him or not? Can I get it or not? How many of you think yes? Yes. It's okay. No? Then he beard yes or no either or get. Tell yes or no da. No.
Yes.
I think yeah. No. He cannot get that 10,000 rupees. The reason is people, she can get it.
What if you promise to pay them?
Correct. He promised. He literally cut one man's kai and he said, I promise. Blood promise. Now, blood inform. Serious promise, intention to create legal relationship. Tell da. Tell da. Yeah, blood to value da. Can I now create or not?
If it promises, yes.
Promise only da. Pinky promise. Now people, remember people. Can I do it? Answer is no. No matter how much of emotion we add, macha, coming and turning off the fire is your duty. I cannot claim it, even though I agreed. It's your duty. Correct. Correct. Very good. Correct. For example, all of you have to clear CA foundation. That's what the rule says. Can you clear it by copying? This is not said in the rule, no. So, macha, whenever you're reading, you have to read as a whole. You have to clear, but not by copying. So you cannot say, sir, offer plus acceptance is there. I will follow only that. You have to follow the entire rule. Here, there is one more rule, no. And always remember, whenever there is general rule, whenever there is specific rule will always prevail over the general rule. This is a general rule. Offer plus acceptance is a general rule. Now, I gave money to Ajmal Kasab, Mumbai attack. Okay. Someone gave money and they said to come and drop one bomb in Delhi. Now someone came and dropped a bomb, offer plus acceptance. Now he's asking for money for doing this job. Should I give it or not? Why? Why the offer plus acceptance? No. But offer plus acceptance, no. Why offer plus acceptance is there? For that, no. For this, you will debate. Exactly. That is, see, your brain is saying, sir, how can bomb become valid? In the same way, it's a law. Law says anything illegal cannot be binding on the parties. In the same way, here it is written, whenever it is your duty, you cannot get a right over it. Meaning you do not have a right to demand money. How can this person go and file a case in the court to claim that money? Correct.
Like only for file that not expected to file that.
Huh.
If the patient thinks that file that,
No, cannot.
duty to perform.
Correct. There also I said the same thing. ಯಾರು doctors family okay. Done now. This is clear, huh? Okay, consideration must be real and not illusory. Magic pro. It should not be lawful, unlawful, immoral, opposed to public policy. Unit 3 will be seeing in detail. Suit by third party or doctrine of privity of contractor. What do you mean by doctrine of privity of contractor? Third party cannot enter into any, he does not have any rights between the parties to the contract. In short, A and B are entering into a contract. C cannot come and poke his nose. Outsider cannot enter into the parties to the contract. Clear? Huh? So if any problem is there, A only should file a case, B only should file a case, not C. That is what they're telling you. Clear? That is only called as what? Doctrine of privity of the contract. But this rule has certain exceptions. The first exception is called in the case of trust. That is, beneficiaries can come and file a case. Any example for a trust? What is a trust? Trust. Hope. Okay, that trust. No, I'm saying organization, institution. Temple trust. Your schools and colleges are a trust. Now, how does this trust work? Someone who has extra money, really good money, he will say, I'm opening one trust. And he will appoint some trustees to take care of that property. Best example, Tata Foundation, Gates Foundation, Reliance Foundation. They have money, they have created trusts. Now, who created it? Ambani created it, Tata created it, Bill Gates created it. And they have appointed trustees to take care of this property. Agreed? Who created it? These people. Who is taking care of it? Certain like board of directors. They are taking care of it. So there is an agreement between those two. Agreed? Same way. Imagine your colleges, your schools. Someone who has created the trust, someone is running the trust. Now imagine if there is a problem in infrastructure. Can you guys go and file a complaint? Can you go and complain, sir? The infrastructure is not good in our college. The building is not right. Can we go and complain? Now they will respond, hey, who are you? The agreement is between me and the trustee. Or the person who created the trust and me. Who are you? Why are you coming and complaining? They are called as beneficiaries. Imagine temples, imagine whatever your religious places are. It is created by someone, it is managed by someone, benefit is taken by you. Can you go and complain? Answer is yes, you can complain. As a beneficiary, you have a right. Hello? Biggest example of Tirumala Tirupati Devasthanam, created by government. One of the biggest trustees we ever had, one of the most powerful person, Vijay Mallya ji, was one of the trustees. Yes, Macha, the TDD trustees, all are like that. I mean, they are all the powerful people only. TDD's trustees. Yes, governors and all are trustees there. Can you imagine? I'm telling you, because fund, நல்ல பணம் இருக்கு. Recently, one case has been invoked. One of the counter. There will be one person who counts, no? So they have filed a case on him saying that he has been taking some money while counting. The counting people will be there. But I hope you guys are understanding what I'm saying. The hundi will be taken, they'll count now. One person has been arrested saying that he has been lobbying some money while counting some money. Now he has made one offer as a compromise. So first thing is he's being arrested, he's been put in jail and all that happened. So the wife and the family said, if at all you arrest him, then we are going to commit a suicide. So they have come for a negotiation. I mean, all of this is happening in trust, whatever I'm saying here. Now, they have offered to pay this fellow, this person, he has offered to pay 26 crores. You imagine now. Now it is left to you what you want to imagine. His salary was 8,000. Nice, no, I've saved. That's how it has become 26 crores. Here, it is an agreement that they have given a proposal to the truster that please do not take any legal action. I will come and give back 26 crores to the trust. So please drop off any legal proceedings. Correct, no? 8,000 per month, 26 crores only, no? 8 3s are 24 plus 2 interest, no? Doesn't work like that. Yeah. So who questioned it? Who are opposing it? Are beneficiaries? Trustee illa. CC cameras. See, the person is caught. She is telling, how did they know, sir? I'm saying. Now, for example, we are beneficiaries. No. Now, for example, what I'm saying is, you also have a right over it. That property also belongs to you. Even though my name is never a part of that agreement, you have a right over it. That is what I'm trying to tell. You will get a right. Understood? Huh? Nice, no? Next one, family settlement agreement. What is family settlement agreement? All any person in our class who has property disputes. Anyone? No, not even one. Surprising. Very lovely. At least one should be there. Much I'm telling you, I'm teaching CA Foundation Law for at least 9 to 10 years. Not even once. I've got a scenario where I asked the same question to the students. Not even once I got a scenario that no one has a dispute. There will be a dispute. And I'll tell you the reason also. You have a dispute? The dispute is anywhere related to the family tree, something like that? Okay. Let us go with one person. 4 generations back. Great-great-grandfather. Great-great-grandfather. Great-great-grandfather had how many grandmothers? Not him. I'm saying in general. Of course, one only. Pati, Patni or what? Now, listen. Law only. Nothing illegal. Now, listen. Hey, don't judge me. Wait. Wait. I tell you why. She's like, my God, disgusting. Wait, I tell you. Even as if it didn't happen. You tell me, and now I'll ask you one question. Very vocal question. You should be okay to accept. Anyone here has more than one grandmother, great grandmother? Hey, same person who said me disgusting. Huh? Yes, sir. Again, second question. I have never received an answer which is none. We always have great grandfathers ki jai. India has the biggest population. How do you think? Now see here, okay. Now see here, people. Now, why litigation is in the deed. Whenever there is a family settlement, what will be happening, people? Generally, whose name will be there? Grandfather, grandmother's name. Grandmother will have some 11 to 15 children. You want me to ask another question? Huh? Your father generation is there. How many brothers and sisters? 11. See, Our grandfathers were the biggest visionaries. Listen, wait, the impact player concept came today. That time only they envisioned. 12 people were there that time only. Today BCCI rules and all. That is the first side vision. Now see here, come back. Now see here, I Bandro. Our age and macha, my grandfather, no. I listen, listen here. I listen, okay, now listen. Now, in the family settlement tree, in the agreements, now the properties, I listen. In the properties, only the grandmother and the 12th person, that is the 12 children's name will be there. Now, what about the brother? After seeing KGF, who is asking who is Raki Bhai. Now, people, Pati, Patni, or Go, it's a valid contract. They also have a right over the property. Now, you take the legal chain. Now, if at all this property has to be sold, you need to get a signature by 1, by 12, plus another 500 people here. No, that's the chain, no? She's saying, how did 500 come? Although QA is done, no? A plus B whole square you put down. You will get the answer. He's asking, sir, prove how 500. Hey, QA class is done, Now you guys only know. A, B, C, D options will be there. Huh? No, correct, no. That's what they're telling you. Got it, huh? Family settlement agreements. Any member of the family. Luckily in India, the family definition looks 7 letters, but there will be 700 people. Yes, no. Now see. So, family settlement agreement, anyone in the family will have a right over the property, whether my name is there or not. That is why machas in India, litigations exist. What happened? Tell me, Kanna. Now she's asking who's the grandfather. Now, that's the reason litigations exist in India. Because you can never get consent from everyone. After 10 years, 15 years, now someone from this family will come and say an objection. Even we had a right, we have not signed. That's how you get a litigation. Whether is it right? Yes, they have a right. Next one, marriage contracts. What is marriage contracts? Any contract made on the marriage, whoever are the beneficiaries of the marriage, they will have a right. Example, people, Khwaja Muhammad versus Husseini Begum. A promised B that if your daughter marries my son, I will give 500 rupees. So the daughter married son and passed away. Daughter ka father passed away. So the daughter-in-law asked that 500 rupees with the father-in-law. You said 500 rupees, you will give it to my father, give it to me only. But the father-in-law said, no. That contract was between me and your father. You are an outsider to this contract. So I'm not bound to pay this money to you. In this case, it was decided marriage contracts for whosoever benefits the contract was made. Even if this person has passed away, the beneficiaries of the marriage can always be entitled for the benefits of the contract. So in this case, the daughter-in-law won the case. Clear? Next one, assignment of a contract. Assignment means what, people? Transfer. I had a right, I gave it to someone. Now they can fight a case. Next one, acknowledgement or estoppel. What do you mean by acknowledgement or estoppel? Acknowledgement or estoppel. What is the estoppel? Stopping someone from changing past statements. Estoppel. Estoppel means what, people? If at all I have made one promise, I cannot go back. That is called as estoppel, right? Yes, I think we had seen one example also. What is the estoppel? Partnership. In by partnership by holding out. Partner by estoppel. You guys would have seen it, right? The same thing applies there. Agreed, huh? Yes or no? Convinced, huh? Any doubts in estoppel or holding out? No? Clear? Okay. Covenant running with the land. What is covenant? Condition. A sold his land to B with the condition that I'm selling you 10 acres. In this 9 acres, you do whatever you want. But 1 acre should always be given back to my son for farming. If a condition is put and sold, you can do anything on the 9 acres, but that condition of 1 acre will always stay with the contract. Now imagine if B sells it to C, the condition passes. I mean, okay. If B sells it to D, the condition will pass along with the sale. So D also can do anything in 9 acres, but D cannot do anything in 1 acre. Clear? Huh? Hello, online you are able to see the audible waterfalls. Joke falls? Online audible ada? Okay, now let's hear. Huh.
Sir, this is valid, sir. Just when you give a restriction, sir. So in the past, they used to sell, but the water is
Which one?
I'm checking the vegetable, but the water you need to pay me.
Huh.
How is that valid?
I didn't get you.
Sir, I'm selling my vegetable.
You're selling your well to me. Okay.
For every bucket of water that you need to pay me.
Ah.
How is that valid, sir?
I mean, why is it coming here?
Sir, because here I'm selling this by complete 90 plus to you.
Ah.
I think that 1 acre I can
No. That 1 acre, you can lease it to me. You can rent it to me, but you're not supposed to demolish it. You're not supposed to build any structure there. So that 1 acre, I'll pay rent. You can lease it to me, but you're not supposed to sell it or build any permanent structure there, because that's the only livelihood they will have. In villages, that's a common place that happens. I will give you my land, but with the condition you have to give it back to me for rent. So they will be in need of money, so they will sell it with the condition that you will give it back to me on lease. They will give you lease, that is the rental amount that will be given. So in your case, that is not the case.
Why does the installer apply in that file?
No, that estoppel is different. See, the estoppel or holding out here means, now why we are telling that, what do you exactly mean by estoppel? Now let us imagine, give me your phone. Give that. Volunteer. Now, nice. CA. Good. Okay. Now, this phone is for sale. I'll sell it for 500 rupees. Who wants to buy? Yes, sir. Okay. You can collect it after the class. Done? Okay. Now, what's your name? No, I said this phone is for sale. Did Nitish say anything? I said it is sale for 500. Did Nitish say anything? Now, when I'm giving it after the class to whoever asked for it for 500, Nitish cannot stop it. Now, this is called as estoppel. When everything was happening right in front of him, he had an opportunity to stop. He did not stop. He does not have a right to stop in the future. Even though it is his product, he will lose the right. Now, why is this coming here? Why is this scenario coming here? Exception. Because who is the owner? Owner is him. But who is entering into a contract? It is me. Now, can he come and stop this contract? The answer is no. He cannot do anything. Now, I got a right, even though I'm not a party to this contract. This is not mine. Agreed? No. See, technically he is the seller. He is the buyer. Then who am I? I get a right here by estoppel. Now he stayed quiet. He has to stay quiet. He doesn't have a choice. This is the estoppel here. Clear? Huh? Okay, last one is contract by agent. We'll be seeing in the agency chapter. We'll be anyways going in detail there. Is clear? Is that clear? Huh? Hello? Okay. Next one, validity of an agreement without consideration, also called as exceptions to quid pro quo. Now, what is that? Quid pro quo means what, people? Something in return. So they should always be giver and taker. That's a generic rule. But this generic rule has certain exceptions. Even if give is there, take is not there, it will still be a valid contract. That is only called as exceptions to quid pro quo. What is that? The first exception is natural love and affection. When will this come into picture? That is what I told you. Now, husband and wife, if they actually want to enter into a contract, when will this happen? Husband wants to transfer a land to his wife's name. Now, can I transfer? Answer is yes. But we saw social and domestic agreements. Tomorrow, husband can come and say, hey, this contract is not valid as per Indian Contract Act. How to prove our intention? They're telling you to prove the intention, you need to satisfy 3 conditions. First one, it should be natural love and affection. It should be parties, it should be near relationship. What do you mean by that? Close relationship. It can be husband, wife, it can be parents, it can be siblings. It cannot be, oh, yes, sir. Grandmother ka friend. Yes, sir. That is not possible. It should be a near relationship. So only then this condition will apply. Agreed? Next one, it must be in writing. Oral will not come into picture. Third one, it has to be registered. If all 3 conditions are satisfied, even if the parties are closely related, you can enter into a contract. Now, this will be an exception to intention to create legal relationship. There we saw on domestic or social agreements. To prove it wrong, you have to follow this. Clear? So if a husband and wife, they enter into an agreement in writing, instrument is registered, then it will be a valid contract. Understood? Hello? Next one, compensation for past voluntary services. Compensation for past voluntary services rendered voluntarily, rendered for promisor. Promisor should be in existence when made. He must have intended to compensate. What is this? What is that? Compensation for past voluntary services. A searched for the, what is that? The wallet. Correct? Now, A went and gave it to B. Now, B people said thank you, and he said, I will give you 500 rupees for coming and giving me this wallet. The moment I made a promise, now I am liable, people. I will have to pay money for this 500. I cannot go back. Now, this is only called as compensation for past voluntary service. Voluntary service is 500. Compensation is me promising to pay for that. I will be liable to pay. What if I have never promised anything? If you have not promised anything, then you are not liable. If you have promised, you are liable. Understood this one? Na? Any doubts here? Na? Illa, not convincing. Allah, you guys understood this or you did not understand? See, what is past voluntary services? Something I did voluntarily. My first thing said what? Consideration will not be valid. If you have done something voluntarily, it must always move on the desire of the promiser. So if I'm doing something voluntarily, it's not a valid consideration. But you did it voluntarily. I promised to compensate you for that. Once I've promised it, it becomes a valid contract. Because I've promised to compensate for that. Then it becomes a valid contract. Understood? Yes. Now, for example, let us imagine someone is drowning in a lake. He went for swimming and he went down. Now he is drowning. Now someone was walking there. Now he gave, now they are all out. Now people, this fellow was having mobile in his pocket. He was wearing a new leather jacket, new shoes. He did not think anything. He went inside. He brought back this person. After bringing back, he's telling, sir, I saved your life, but I lost my mobile. I lost my leather jacket. Can you please compensate me for this? Now you tell me, is this person liable to compensate? Is he liable? Not even 1 rupee. Because same thing, first condition what? Consideration must always move on the desire of the promisor. Did I ask is what I will say. Even though it will be inhuman, yes, I am not liable to pay even 1 rupee. But imagine after coming up, I said, thank you so much for saving my life. I will give you 20,000 rupees for saving my life. It becomes a binding contract. Are you getting the point? Now for this 20,000, am I doing something else again? No, no. You are giving 20,000. What am I doing now? Nothing, no. But why am I getting this 20,000? For whatever I've already done. That's what is called compensation for past voluntary service. Is for 20,000, am I getting something in return now? No. Something I'm not getting now, no. Yes or no? That's why it's an exception. Clear, huh? Yes, sir. Okay. Next one, promise to pay a time bar debt. What do you mean by time bar debt? So if A has taken loan from B and A did not repay, B people should go to court and file a case. Within how many days? B should go and file a case within 3 years. It is written in the act that you have to go and file a case within 3 years. If I do not go within 3 years, people, I will lose a right to go after that. Now let us imagine 3 years is done. We took loan in 2020. The 3 years was done in 2024. The contract is done. Now can B go and file a case now in the court? Answer is no. B will lose the right. But A is really good fellow. A came and said, B, I will still give you money. I will write one more check in 2025. I'm so sorry I could not pay. Then now I have money. I'll give you money within next 1 year. I will freshly sign one more agreement. So A signed one more agreement. Imagine like a promissory note saying that I will give you money next 1 year. So there is a second agreement coming into picture. Me telling again I will pay money. Now tell me, for the second agreement, what did B give again? First agreement, you gave money, I agreed to repay back. Give and take is there. For the second agreement, I am agreeing to repay it. But what have you given? Have you given something? No. So a person agreeing to pay a time bar debt, it need not have give and take. It will be for the same thing, whatever I've taken 5 years back. That only I'm agreeing to give it back. For this, a quid pro quo need not exist. Give and take need not exist. That's the meaning. Understood? Agreed? So now I'm agreeing to give. What am I getting again? In return, nothing I'm getting, no? But it is still valid. That's why it's an exception. Clear? Next one, to create agency. When we are seeing agency chapter, I'll tell you. Gift, of course, it's an whenever someone is gifting you, what will you give them? Nothing. That's why it's an exception. Bailment. What will you give in return? You take your friend's notes to copy. What will you give in return? Chocolate. You charge it, rent and all is there? No, no, free only, no. You're not charged. Then is it a valid contract? Answer is yes. When you're seeing bailment, we'll see. Charity. Charity. Charity is a valid contract. Is charity a valid contract? People remember, yeah. Okay. There was one patient who is suffering from cancer. You know this, they do this fundraising, no? So A messaged, A got a message that we are raising funds and all. A said, okay, I will contribute 10,000 rupees. That time people, they had not collected any money. Even 1 rupee is also not collected. A said, I will give you 10,000 rupees. But I need 25 days time because I am waiting for my salary. So the hospital people or the charity people said, okay, sir, we don't mind. Now, after 25 days, people, he checked what is the amount collected. They have collected people around 1 crore rupees. Now, meanwhile, what the charity people have done, because they got a net amount. They have put the total, how much we are receiving. They had money. They have started the treatment for the cancer. Now, what did A do? A saw the total amount they have collected. That is 1 crore. Now, A thought, hey, I promised when you guys did not have any money. Now you guys have money. I have not yet given. I have given a word. I promised that I will give. When you guys did not have anything. Now you have everything. So A wants to take back his promise. Now the charity house is saying, no, how can you take it back? No, you have to give us at any cost. They have come to you for your opinion. Now you tell me, can A take back his promise, or A should give this charity amount? A should give. A should give, or A can take back? Charity. A asked one thing, hey, I am giving 10,000. What am I getting in return? Charity. Is not liable? Not liable? Correct. Obligation. People remember the exam question, people, provided if the charity people have incurred any obligation, treatment has started, treatment has started, 10,000 becomes an obligation. You will have to pay. Scenario number 1, treatment started. A will have to pay 10,000. I cannot take back because the charity house has created some obligation for this 10,000. Keeping your money also in mind, they might have planned something. You cannot take back your money. Scenario number 2, operation not yet started, obligation not yet started. A can't take back money because it's a charity. You cannot enforce it. And obligation also is not started. Obligation means what? Operation not started. So there is no fixed payment that these people need to make. In such case, A can take back money if no obligation. A cannot take back money if there is any obligation. Exam question, remember, important. Clear? Case law quoted. Kedarnath versus Gori Mohammed. Same case law. If any obligations have been taken up, a charity amount cannot be cancelled. If no obligation is taken up, then charity amount can be cancelled. Kedarnath versus Gori Mohammed. Is clear, all of you? Hello? Pakka? Done? Okay. If you guys want, you can take some 10 minutes break. You can quickly come back. We'll again continue. Probably class can go up to 1:15. That's all. Okay. The next unit, unit 3, people, other essential elements of a contract. Capacity to contract, section 11. Okay, let us start with the first one, other essential elements of valid contract. Now we are coming to the capacity of parties. The first one is called, people, you should have been major. So what are the rules regarding the minority? Is the minor, hello? Yes. Is the minor liable for any terms of the contract? Is a minor liable? Answer is no. A minor will not be liable for any terms of the contract. Only exception is if it is for necessities like education, shelter, food, and not only that, remember, if there is any dependent for the minor. For example, there was a minor whose age was, let us imagine, 16-year-old. He had a grandmother, probably aged 82. There was a neighbor who gave money for the minor's education and also gave money for the medical or any expense of the grandmother. Remember, for whatever the assets the minor has, the minor will be liable both for the education money, whatever he has taken, and also for the dependent, whatever money has been paid. If there is any dependent on the minor, if there is a money given for that, even for that also minor will be liable. So if the money is, say, for education, if it is coming to 1 lakh, if the medical of the grandmother is coming to, say, 2 lakh, the minor's assets will be liable for the 3 lakh. So you are liable for the money given to you, also for the dependence on you. For both, you will be liable. When I say you, it will be your assets and not personal liability. That means what? Sir, minor has zero money. Will minor be liable? Answer is no. Sir, minor has a land worth 2 lakhs, but the liability is 3 lakh. The minor will be liable to the extent of 2 lakh only. So how much ever is your assets, to that extent you are liable, not beyond that. Clear? Yes, sir. Okay, that's what they're telling you. The rules regarding minor agreements. First one is it's a void contract. It's void from the beginning. Sorry, void agreement. It's void from the beginning. It's void ab initio. Case law Mahari Bibi versus Dharmodas Ghosh. A minor agreement can never be ratified. Meaning, when he was 16, he has taken loan. When he is 18, you cannot make it a valid agreement. You cannot tell him to be liable for whatever he has taken while he was 16. You cannot tell him to write one more agreement while he is 18 to pay all the debts he took it while he was 16. Such things cannot happen for a minor agreement. Here, so minor agreement can never be ratified. Ratified means you cannot make it valid in the future. So imagine if I have taken a loan at 16, technically void ab initio. I'll call him after he becomes a major. I tell him, hey, you remember you have taken loan when you're a minor. Now that you promise to repay now, even if he signs, it will not bind him. There is only one exception for minors ratification. It will come in partnership. When it comes, I'll tell you. But remember, clear? Okay, next one. He can be a beneficiary. Can he be a beneficiary? Answer is yes, he can be a beneficiary. That is, partnership is the biggest example. You can be eligible for the benefits, but not for liability. Can he plead minority? Answer is yes. That is, he can go and tell any day, I'm not liable because I'm a minor, so I'm not liable to repay any loan to you. Can I go and tell it any day? Answer is yes, I can go and tell it. Next one is, his estate is liable for necessaries, which we saw. That is, you are liable for the education and for all of that, your estate. Estate here is your property. The property will be liable. He enter into contract by guardian, meaning, can he be a shareholder? A minor cannot be a shareholder, but if he wants to do it, a guardian can enter into a contract on his behalf. The best example is your school education. Who signed it? Parents signed it, and that's what is called as guardian. So you cannot enter into a contract. You can, if you want to enter into a contract, it has to be through your guardians. Clear up? Hello? A minor can never become insolvent. Why? Because he is never liable for a contract. Then how can he become an insolvent? When you become insolvent? I've taken more debt. I'm not liable only. So how can I become insolvent? A minor can never become insolvent. You can never demand specific performance against the minor. I'll tell you what is specific performance when we are doing breach of contract and its remedies. There I'll tell you. Can be an agent. A minor can be an agent. We will be seeing this in more in agency chapter. You cannot bind your parent or guardian. They have asked once or twice a question in this point. A minor cannot enter into a contract and say, my parents will come and pay the money. If the other party believes on that and enters into a contract, still the parents are not liable. A parent can never be bound by a minor's agreement. Now, for example, imagine you come and sit and you say, sir, our parent will come and pay tomorrow. I cannot hold your parents liable for whatever agreements you guys made on their name. Clear? Hello? If there is a joint contractor, what do you mean by a joint contract? Imagine a major and a minor have borrowed money. Minor will not be liable. Major will be liable for the entire money. Together we borrowed 2 lakhs. In that 1 lakh is taken by major, 1 lakh is taken by minor. But together we have to repay 2 lakh. But who will repay? Major's liability will always be there to repay 2 lakh. Next one is surety will be liable. What do you mean by that? Sir, minor borrowed 2 lakh rupees. This contract was given a surety by a person called B, who is a major. Minor is not liable to repay, but surety, if he is a major, he will have to repay. He will be liable for the contract. Minor, can he be a shareholder? Directly, No, but can be represented by guardian. He is liable for torts. What do you mean by tort? Tort means civil wrong. If you abuse someone, if you hit someone, if you do trespassing, for all of this, you are liable. Of course, because tort is a civil wrong. That's why it is coming under breach of contract. But are you liable for any murders you do? Is a minor liable? Can he be arrested? He will be arrested, but the treatment will be different. You will not be punished, but you will be put in school, juvenile board. Yeah, that is education will be given to you. You will not be punished, even if it's a what is that? A murder. The example for that is your master movie. That is what Vijay Sethupathi does. No loophole. The murders will be done by the minors because they will not be punished. Yes. Yes. Tort is a civil wrong. Criminal law, minor will be liable. Clear? Okay, sound mind. What is sound mind? A person entering into a contract should be of a sound mind and not a unsound mind. What do you mean by unsound mind? A person who is insane. That, but remember, if a person is temporarily capacity not correct. So a person who is temporarily unsound, but generally sound mind can enter into a contract when he is sound. For example, from morning to night.
Sir,
6 hours. From morning to night, he is sound mind. From night, he becomes little tight. When Atma meets Paramatma. Yes, sir. Can you understand? Oh, yes, sir. That is when I'll be with full clarity. So, whenever intoxication happens, you are an unsound mind person. You are not eligible to enter into a contract. So whenever you are unsound mind, you cannot enter into a contract, but sound mind, you can enter into a contract. The same way applies to other person also. A person who is usually unsound, but temporarily sound mind, can enter into a contract when they are of sound mind. Who is that person who is usually of unsound mind? Generally, people, those nowadays it's not something new, right? A lot of clinics who deals with the depression, all those ADHDs, your border personality disorders, not something new, right? I hope you guys would have all heard of it. Depression, so I need not explain it to your generation at all. If someone is going in the road, I'll say, why da? Sir, depression. No. For why only depression? No? Yeah. So that is what? That is called an unsound mind only, no? Borderline personality disorders. Unsound mind only, no? ADHD, so many things are there, no? No? New schemes, sorry, scheme Allah, no? New things and all are there now. And the person should not be expressly disqualified. Who are expressly disqualified? Foreign sovereigns and ambassadors. This is not card of Machan. Ambassador here is nothing but the people representing foreign governments. Why? That is, why are we disqualifying them? So that you guys do not mess up our relationship with them. Imagine Trump comes here. You enter into a contract and you cheat him. He will already he is taking revenge on the world. He will take more revenge. So to not spoil the cordial relationships, we disqualify them. If you still want to do it, you can do it with central government's approval. Yes, sir. Next one, alien enemy, Shoaib Akhtar, insolvent, Vijay Mallya, convict, Sanjay Datta. Correct, no? All these people cannot enter into a contract. Convict, correct, no? Convict is what? A person arrested. Deboss. Darshan can enter into a contract? No? Darshan can enter into a contract? Yes. Darshan can enter into. Darshan is an accused, not convict. Sanju Dada was convict. Convict is case filed proven. Now Salman Khan, you were telling me that time. Salman Khan was accused. There was some case on Salman Khan. No? Yes, no? What is the case? He drove over people. Is it true? Silence. Meditation. Correct? No, we don't know. I mean, he did not do it. He's out free. That means he has not done it. So when a case was filed, that means he was an accused. Sanjay Dutt, there were some allegations of a lot of things, but the case was proven. He was proven guilty. He was in jail. He was doing labor. He was doing carpentry work. 40 rupees per day was his wage. Yes. Sanjay Dutt was a convict. When he is in jail, he cannot enter into contracts. Now, people generally ask, sir, what if they are released? Then how did KGF happen now? KGF will villain now. When did it happen? After him coming from jail only now. Then convict is only as long as you are in jail. After that, you are a free man. You can do anything. Corporations is nothing but people, companies. This is nothing but people, MOA, nothing but people, ultra wires transaction. So your object clause, whatever is given, you are only supposed to do that. You're not supposed to go beyond that. If you go beyond that, it is considered as disqualified. Clear? Next one, people, free consent. The first one under that is called as people coercion. The next essential element of valid contract is nothing but free consent, meaning no one should have forced you to enter into a contract. Coercion is nothing but people force. What is the difference between undue influence and coercion, people? Coercion is nothing but which focuses on something which is punishable under your BNS, not IPC, BNS now. So if you have done something punishable there, murder, threatening to kidnap, now for this you will be imprisoned. If you have done something like that, that will come under coercion. Sir, undue influence. Hey, if you don't give me your mobile, I'll put 5 months less for you. That this and all is threatening. If you do not give your mobile, I'll not allow you for tomorrow's class. Probably as a student, you might be worried, but is it something like life and death saving decisions? No. For this, should I be punished? Say no, da. Silence. Yes, for this I need not be punished, but what I did is wrong. For this, I need not go and sit in jail and all. That's what is undue influence. The nature of offense will be less. And there is always a relationship between the parties, like teacher, student, doctor, patient, debtor, creditor, master, servant, employer, employee. There is always a relationship. And there will always be one party in a higher authority, one party in a lower authority. So one person, if he misuses his dominance, it is called as undue influence. Clear? Yes, sir. Uh, See this question? I mean, I'll take the next question also. This we should have seen it before only. Mr. A was running an orphanage. His friend Mr. S, a philanthropist, agreed to donate 2 lakh for the treatment of a child who was suffering from cancer. In an emergency, Mr. A incurred 1.5 lakh on the treatment of the child. Now, Mr. S refused to pay. Whether A can claim 1.5 lakh from S with reference to the provision of Indian Contract Act 1872. Can he? What grounds? Charity will become a debt if at all any liability is undertaken. Example, I will write Kedarnath versus Gauri Mohammed. Clear? Huh? Okay. Okay, see this question. Chandan was suffering from some. Now I will do see. Yeah. Chandan was suffering from some disease and was in great pain. He went to Dr. Junjunwala, whose consultation fee was 300. The doctor agreed to treat him, but on the condition that Chandan had to sign a promissory note of 5,000 rupees payable to the doctor. Chandan signed the promissory note and gave it to the doctor. On recovering from the disease, Chandan refused to honor the promissory note. State with reasons can doctor recover the amount of promissory note under the provisions of Indian Contract Act 1872. Why? Huh? It is our duty to perform. Okay. It can be, that's why I'm saying it will come under both. You can say that it is a legal duty to perform. Correct. Now, you do not know how much of it is legal duty. How much of it is legal duty? He's saying I'm charging 5,000 as fees. What if that itself is his charges? So, you got the point? Why you guys are getting confused? In the example which I told you, I clearly told, sir, 5 lakh is my fees. You have to pay me extra 5 lakh if you survive. Surviving is your fees. I mean, surviving is your duty. For that, you are not supposed to charge extra. Are you getting the point? Here, what are they given? 300 is my fees. But for the same treatment, nothing, surviving and all, nothing is there. But for that, I'm charging 5,000. Where does this come under? What is the answer? Performance of? What one is legally bound to perform? Okay, under that, can I recover or no? No. Remember, people, the answer comes under undue influence, mental distress. There is a specific point under undue influence. A doctor and patient shares a bond. Doctor is in a dominant position. Now I know that this treatment is essential for the patient. Using that, if I'm charging more fees, it will come under undue influence, under the exact topic called as mental distress. You guys remember seeing something like that? See, that's where I tell you, don't go generally. If there is a specific point where you need to remember, there will be a specific point. Understood the complication of law? That's why I told you, focus on Companies Act. Yeah? Now come see. An undue influence can be used against a person to get his consent on a contract where the mental capacity of the person is temporarily or permanently affected by the reason of illness or. Now, because of that, what has happened? There is a person whose treatment generally he charges 300 rupees. But the doctor says, for your treatment, you sign me a promissory note of 5,000 rupees and give it to me. I'm charging more. After getting cured, the doctor asked him to pay 5,000 rupees. Now the question is the patient liable to pay this 5,000? Answer is no. I'm liable to pay your fees. How much ever is your legal fees? For that much I'm liable. Anything beyond that, I'm not liable because you misused your position. Now you know that I will pay. I have to pay. You're misusing that. Sir, to understand it better, tell us. Now imagine people, you go to a hospital today. You say that there is a little leg pain. Now they will tell people, go for an MRI, go for an X-ray. Now why? If you can prove it is a misuse of power, you will come under this scenario. Because there is a doctor, there is a patient. If they can prove, no, for your treatment, all that is required, if they can prove, then no, they will not be liable. If you can prove for your treatment, all that is not required, then you will win. If they can prove it is all required, they will win. Understood? Exam question. That's why I put it under tricky question. Are you getting? Wherever people have chosen this over that, those questions only have taken. I told you that firefighter example also. People have chosen the other one. Past voluntary services, compensation to pay for past voluntary services. People have written answer that term. Getting the point? Hello? See. Undue influencer. From the facts, Chandan signed the promissory note under undue influence applied by the doctor. Hence, Junjunwala cannot recover the amount of promissory note but can claim his normal fees from Chandan. Agreed? Huh? I hope you guys are understanding. So, when and all can this scenario exist? When and all undue influence can exist? Undue influence can also exist. One of the other Exam question they have given us. Now say for example, a father enters into a contract with his son. Of course, both are majors. A father agrees to sell a certain property of his to the son for almost 50% more than the market price. The son agrees to buy, but later son realizes that the price that the father has offered to the son is almost 50% more than the market price. The son now wants to cancel the contract. Can the son cancel the contract? Under what will it come? Undue influence under which condition? You know, undue influence has more conditions. One I showed you is mental distress. Where will this come under? Which one? Fiduciary relationship. Fiduciary is what? A relationship of trust. A son will believe in the father. So son believes in the father that a father would never cheat me. On that trust, I would have entered into an agreement. And now if father is cheating you, you can go under undue influence only, 100%. If you can choose the right sub point, that's the best. I will write under fiduciary capacity. Understood? I'll give you one more example. There is a farmer who is in dire need of money. You know, right? You literally look at our movies and all, you will know. There will be that farmer who has nothing, he will be very lean. They will show the movie like that only. So, and that scenario, we will go to the, what is that? The zamindar of that particular village. He'll go and ask for money. What will the zamindar do? You want, I will give you. What do you have? I have gold. I have property. Then do one thing. Give me your land documents. He take the land documents and I'll give you the loan at a rate of interest of 4% per month. That is like 48% per annum. The bank interest will be around 15% per annum maximum. Now the farmer takes the loan, but while repaying, the farmer is going to the court and asking for the help that I will not repay 48%. Now the question is, can the farmer negotiate, renegotiate, or can he cancel this contract? Is it possible? Under what grounds? Unconscionable bargains. What is unconscionable bargain? The creditor knows the scenario of the debtor and I try to misuse my capacity. See, I know you don't have a way out. You need money. Because of that, I'm charging higher rate of interest on you. In such case, I can go to court. I can get the rate of interest revised, allowed. If I go to court in this case, what happened? They will say the loan agreement will be valid, but the rate of interest has to be reduced. You charge 20%, that's okay. I'm not saying you have to charge 15 only. You charge 20, it's okay, but it should not be unreasonably high. It comes under unconscionable bargain, meaning non-reasonable bargain. Bargain means always debtor, creditor should come. Hello?
Yes.
Pakka na? Sure. An employee has a wonderful bike. The employer forces the employee to sell the bike. If not, he said, I will not give you the promotion this year. Employee sold the bike to the employer. Can the employee cancel this contract? If yes, what is the ground?
Fiduciary position.
Real and apparent authority. What do you mean real and apparent? Real and apparent. Apparent. The word apparent means people. By looking at the face of it, anyone can say employer, employee, employer in the dominant position. Real and apparent means that. Apparent means on the face of it, it is visible that one person is in a dominant position. If the person in a dominant position is taking the advantage, then in such case, yes, you can go and cancel the contract. So I gave examples for all four. Real and apparent, meaning on the face of it, it is visible. Fiduciary relationship, nothing but a relationship which is involving trust. Example, you and your bank shares fiduciary relationship, matter of trust. All your bank accounts, your money details, everything is with your bank. On what basis you guys have given? On the basis of trust. What if they give it away to someone? What if your OTP is shared to someone? Understood? Next one is unconscionable bargain, debtor and creditor, mental distress. It happens only in the case of doctor and patient. So if doctor patient comes, the first thought that should come to you is there is this one. First is undue influence. Under that you need to think of mental distress. That is how you need to dissect. Getting the point? Yes? Hello? Understood? Okay. Unconscionable bargains. Okay. Undue influence, I hope this is clear. Dominating position. Okay. Next one is fraud. What is fraud? A person who is knowingly, a person knows that what I'm saying is false, but still I will say it is true. Meaning what? This pen, while I was outside, it fell from my hand. It did not write. I know it is not working, but I'll still come to the class and say, people, it's a very finely working pen. I know it is not working, but I'll say it is working pen. Now, what I did is called as fraud. What is my misrepresentation? Now, I kept it here and I went for a break. While I went for a break, someone had dropped this pen and has clearly kept it back. Now, I came back and said, people, this is a working pen. Now, do I know that it's not working? I have zero clue over it. Now, this is called as what? Misrepresentation. That's the difference. In fraud, people, you know that it is wrong, but still you say it is right. In misrepresentation, I don't know it is wrong. That's why I say it is right. That's misrepresentation. Is it clear? Now, let us imagine this pen is not working. I know it, but I'll come and say, people, this pen is for sale. This pen is not working. I know it, but I will not disclose. I will say this pen is for sale. Now, say for example, Nitish purchased it. After going home, he saw that this pen is not writing. Now, he is filing a case on me that it's a fraud. Tell me, is it a fraud? Understood the question? This pen is not working. I know. I still sell it to Nitish. Nitish pays money, takes home, writes and practices. It is not working. He wants to file a case on me. He's saying what it is a fraud. Is it a fraud? Is it a fraud? Why? Because knowingly I sold it. Agreed? Yes, sir. What I did is not a fraud. There is something called as KVA tempter. You guys would have studied also, no? Mere silence is not fraud. I did not disclose. There no one in the world will disclose their loopholes. Understood? Is it a fraud? Answer is no, not under the law. If the defect is, it's simple. He is trying. Now people tell me, when you are buying a 10 rupees pen in a stationery shop, what is the first thing you guys will do? Remove the cap or sign. Correct? On 10 rupees, why did you want to sign? You take home directly now. Why did you do that sign? Checking. KVA tempter. Let the buyer be aware. So, whatever. Now, don't you think he can just he can come and do this? Now, did he do that? So, remember, if the mistakes was unidentifiable, meaning with bare eyes you cannot find it, with reasonable care you cannot find it, then what I did is a fraud. Now, how do I tell it, sir? Let us imagine that I'm selling you this furniture. Inside this table, there is a crack. Now, if it is visible for you. What do? I cover it with this laminate. Now, the crack is inside. See, how will anyone test? They will check, okay, everything is correct. What, he will stand on this and he'll jump? No one will check it like that. Now, after some 5-6 days, it will break. Now, whatever I did, is it a fraud? Answer is yes, because I hid my mistakes. In the previous case, I did not hide it. If you had checked it, you would have made it out. That's the difference. So, whenever the mistake is evident, if you check it, if you can find it, and if you did not put your effort, seller will not be liable. Seller by default is not liable to disclose the mistakes. He will not disclose. It is not a fraud. Unless and until it is a contract of Uberima Fidus. What is that? Contract of utmost good faith. What are the contracts of utmost good faith? Your share allotment contracts, prospectus, IPO. If you do not disclose even one letter, whether intentional or unintentional, it is fraud. Insurance contracts, everything is a fraud, whether you disclose or you don't disclose. Marriage contracts, by default is fraud. If you do not disclose. Marriage contract, see, why is marriage contract coming here? What if a person had a financial burden, lot of debts, did not disclose? What if a person had health issues, did not disclose? I only know one case where, the boy had one of the medical issue that was not disclosed at the time of wedding. But after 2 months, they figured out that there was generally it was a problem of, fits. The fits problem was there. The girl's family filed a divorce application and it went through with maintenance because it was a cheating. Now, the boy could have also said, no, you should have asked for it. Correct. Who will come and check that marriage? You have any health issues? BP, sugar? I don't know. He's like, I don't know, sir. Kya beta? So that's why it's an exception. See, exception meaning even mere silence will be a fraud. In a insurance contract, marriage contract, in a prospectus, it will be a fraud. Clear? Hello? Pakka? I hope this is clear. Fraud. Next one is misrepresentation. What is misrepresentation? False, true, false. Understood? What is misrepresentation? Even I don't know that there is a mistake in the product I am selling. Yes. In such case, what will I tell it as? I will call it as mistake. Misrepresentation. Fraud is something I am aware of. Misrepresentation is something I am not aware of. Simple? Hello? Okay. Only difference between misrepresentation and fraud is people. One is that you are aware of. In misrepresentation, you will not get damages. In fraud, you will get damages. Because you did it intentionally. Compensation, you will get it. In misrepresentation, you will not get damages. What do I mean by that? Let us imagine I sold this pen under fraud, under misrepresentation. So, if at all I sold it under misrepresentation, if the value of the pen is 10,000, he can give me back the pen, I'll give him back the 10,000. If it was sold under fraud, he will give me back the pen. I will give him 10,000 plus some extra money for cheating. Clear? Yes, sir. Okay, last one is mistake. What is mistake? By mistake. Mistake of law or mistake of fact. What do you mean by mistake of fact? What is mistake of fact? Generally, it happens in Arivu, mistake of fact. Okay, I'll not take that. I'll take one other example. Okay. No controversies. Okay. Now, say for example, I go to a okay, easiest one. I order something on Amazon. What do I order? Let us imagine I have ordered for a shirt. But Amazon has sent me some other product. It can be same shirt, but of a different color. It can be a different product. I have ordered for a shirt. Probably I got pants. And I believe such thing definitely would have happened with you. Kadanto, it might have happened. Different product. You have in a return item only. You have that option. No, you received a different product. You have that option. Yes. No, sir. This is called as what? Mistake of fact. I have ordered for shirt, but what you sent me is pant. Now this is only called as what? Unilateral mistake. Why? I know what I have entered into. I want shirt only. But you are under a mistake. One party is under a mistake. That is called unilateral. Unilateral mistake will always be valid. If it is a bilateral mistake, it is considered as void. What do you mean by bilateral mistake? Both the parties are under a mistake. Now, for example, A said, I want to sell my car to B. B asked how much. A said, I will quote 5 lakh. B is like people, A always uses BMW. He is like, my God, that car is selling for 5 lakh. B said, okay, I'm okay with it. When should I come and collect the car? A said, come and collect tomorrow. Now, people, B came tomorrow. So, B Papa went in proper formals and all, oh, nice car and all. So, he came and asked for keys. He gave. He said, why this keys? He said, this is the car I'm selling. Where is the car? It is standing right in front of the home. Which car? Probably Nano. Tata Nano was standing. There, that car you are selling, huh? That car only. Which car you thought? I thought you are selling your BMW. People, this is called as what? Bilateral mistake. I thought you are selling BMW. He thought he's selling Nano. I am thinking it is a everyday car you are using. Who knew that you had one more car? This can come under two things. This can be vague also. It can come there also. Consensus ad item, meeting of minds. It can come under offer, vague. It can be under consensus ad item. Remember, bilateral mistake is nothing but absence of consensus ad item only. Bilateral mistake. You are also under a mistake. I am also under a mistake. So this is only called as what people mistake of fact. What do you mean mistake of law? Mistake of law, people, it depends whether it is an Indian law or it's a foreign law. If it's an Indian law, people, you cannot treat the contract as void. The contract will be valid only. Example of Indian mistake, people, mistake of Indian law. Imagine you get into a train. As per Indian railway rules, you have to buy a ticket. You cannot say that I was not aware. Even if you say you're not aware, you will not be left. They will not say, okay, get down. It is considered as a valid contract. You have to buy a ticket. You did not buy. You have to pay damages. It's considered as a valid contract. Mistake of Indian law. What is considered as mistake of foreign law? Mistake of foreign law is you do not know. Now, for example, people, recently that MDH Masala company, there was an issue on MDH Masala company. What happened? They sold certain masala products to Australia. See here, MDH and Everest, Indian spices face heat over global rejection. MDH spices were rejected due to the presence of bacteria, something. Some and all content is there. If we go in detail, you'll get there is some element which is used more than a prescribed limit. So in these countries, that chemical cannot be used. They are not like Indians. We can digest fertilizers also. They are sensitive people. Yeah. So no, they said that those elements cannot be used. Now in India, it is valid. MDH Papa, like that only they thought they are also insensitive people. They sold. But when they received the first sample, when they did a lab report, it came out that there is a particular chemical beyond what is prescribed limits. Now, you imagine the consignment, almost some crores, hundreds of crores worth of consignment was sent. Now, what will happen to that? Who will bear the risk? Seller thinks it is valid because in India it is valid. Buyer thinks it is valid. He thinks it is not there. I did not know that is restricted there. Now, in such case, what do? We come and treat a mistake of law as mistake of fact. What do you mean by that? If one party knew it, then you will treat it as valid contract. If both of them did not know, then it has to be treated as a void contract. It becomes void. You have to return back the money. You have to take back the goods. If one party was aware and still you did it, it is a valid contract. Then breach of contract will happen. Damages and all will come into picture. That's the meaning of mistake of foreign law is treated as mistake of fact. That means unilateral, valid. Bilateral, void. Is this clear? Yes, sir. Hello. Okay, next one, legality of object and consideration. Forbidden by law. What is forbidden by law? You cannot do anything which is forbidden by law, like child marriage, smuggling, and all that. Defeats the provision of law, meaning if any law has clearly given one right, you cannot take away that right. For example, minor agreement is void. You cannot say that condition will not apply to my contract. Such condition will become void. Next one, fraudulent smuggling and all. Involves injury to a person or a property, like threatening, damaging someone's property. If at all a contract is made for all of that, it will be considered as unlawful object and consideration. Immoral, what is immoral? Immoral, there is nothing called as legal or illegal. Now, for example, the marriage I told you, it becomes immoral. It's not legal or illegal. It's immoral. Correct, no? Now, for example, there was again a case. A and B are a married couple. C has told B, you divorce your husband, I'll give you a compensation of around 1 crore and then you marry me. There was an offer made by one of the party and B has taken up the offer. A real life case. Now, is it legal? Is it legal? C gave an offer to B to divorce A and come and marry him. Is it legal? Is it written somewhere? This is neither legal, neither illegal. Nowhere it is written. It comes under immoral. So such contracts will come under unlawful object and unlawful consideration is what they are telling you. Understand the difference between legal and immoral. Illegal is somewhere specifically written, you cannot do it. Clear? Okay. Consideration opposed to public policy. So if at all you are entering into a contract, but that particular thing is opposed to public policy, such things are considered as unlawful. What is it opposed to public policy? First one, trading with enemy. Your TikTok, PUBG, alien enemy, Shoaib Akhtar, everything will come there. It is considered as unlawful because it is not good for the public. Next one, trafficking of public offices and titles. What is trafficking? Trafficking means people nothing but selling. Public offices means what? Government office. You want to become what? Commissioner, huh? I'll tell you 20 lakh rupees it will cost. If I say that, that means what? You're selling a public post, public office, a designation. It is coming under this. It is considered as opposed to public policy. Titles is what? Padma Bhushan, Padma Vibhushan. I'll tell you, give me 1 crore, I'll give you the title. Understood? Huh? Yes, sir. Next one, agreement creating monopoly. Airtel and Jio will come and say, this is the tariff. What will you do? Your monthly package will cost 1,000 rupees. Both will charge the same thing. Do you have other go? Huh? That is called as creating monopoly. Any agreement creating monopoly will always defeat or it will have a very impact on a public. That's why it is coming under public policy. Considerations opposed to public policy. It is not in the welfare of the public. They will suffer. Understood? Huh? Okay. Next one. Marriage brokerage agreements. Long back it used to happen, people. There used to be brokers who used to do liaison business. Meaning what? A and B. They will go and tell, hey, you know, A, wow, full assets. They have full property and all. Very nice. You go marry. No, why are they doing it? Because they get commission. Such agreements are considered as invalid. Remember exam-based question. Are Naukri.com, marriage brokerage, whatever, bureau, matrimonial sites, are these valid? Answer is yes, they are valid because It is just a website which gives you an information. They are not doing any business of convincing people. They will just give you the data. For that you are paying. And that's why it is not coming under this objection. It is not opposed to public policy. I hope you understand the difference. So your matrimonial sites, they will charge you money and they give you access to the website for 1 month. You can shortlist the profiles and you can personally contact. They are not doing anything between you guys. But marriage brokerage agreements here are nothing but a person, convincing you for the purpose of commission. They say, no, no, you have to get married. That is illegal. Yeah. Okay. Next one. Interest against obligation. What is interest against obligation? Interest against obligation. Imagine people, government offices done. They need to buy some products from us. They have to buy from, probably let us imagine a government wants to buy some stationery items. If government wants to buy anything, people, they have to buy it in a tender, bidding. Now, the government officer, there is 3 proposals. One proposal is 10 rupee per kg, 20 rupee per kg, 30 rupee per kg. This 30 rupee per kg person said the officer, Macha, if you give me the contract, I'll give you a commission of 10 rupees. The government officer's job is to what? Is to select the bid whichever is most beneficial to the government. So he should have selected 10. But what will the government officer select? 30. This is only called as what? Creating an interest against obligation. Your obligation is to select 10. You're creating an interest for 30 because you're getting 10 rupees. Such contracts are opposed to public policy. Clear? Hello? Consideration unlawful in part. It can be severed, then such part shall be valid. What do you mean by that? A enters into a contract with B. I want your land for lease. I want to cultivate some crops. B gives the land to A. Now, is this contract valid? On the face of it, yes. Now, what did A cultivate? On the first part, he cultivated rice, paddy. Second part, he cultivated A. Yes, sir. What did he cultivate? Second part. Something is there. One dosha irukku. They are dropping every bottle possible there. So, in first part, they have cultivated rice. Second part, yes, sir. I don't know what is that. They said, I don't know what is weed. Yes, sir. Now, people, you tell me, is it a valid contract? Can I say the entire contract is invalid? Unlawful in part, this will be invalid. Lawful in part, this will be valid. Simple? Yes, that is what they're telling you. Next one, people, stifling of prosecution. What do you mean by stifle, people? Stop. What do you mean by that? You cannot make a trade of felony. Felony means what? Crime. Yes, sir. Felony means crime. You cannot make a trade of felony, meaning you cannot make a trade of crime. If a crime has taken place, you cannot settle it. You have to go to court. That's the meaning of you cannot stop the prosecution. Prosecution means what? The formal procedure, court procedure. You cannot stop it. Imagine A killed B. And A is telling, I will offer some compensation to the family. Don't come and file a case. Don't come to the court. Don't come. Witness, I'm telling you, don't come to the court. Such things you're not supposed to do. That is the meaning of stifling of prosecution. Opposed to public policy. Clear? Next one, maintenance and champerty. What do you mean by maintenance and champerty? A and B. Let us imagine. B has okay, let us imagine A has taken some land from B by force. A has taken some land from B by force. That is coercion, can I say? But A has taken land from B by force, but B does not have that strength to go and fight this case in the court. He doesn't have money, he doesn't have guidance, nothing. So C comes and says, you do one thing, I will give you money. You go and fight this case in the court. Now B is asking, what do you want in return? If B asks, whatever I gave you, give me back the same thing. Or once you win the case, you do one thing, you give me 2% of whatever you win. Now, whatever C did, the helper, that is only called as maintenance and champerty. When someone is helping you financially to fight your case, in return, they may expect their own money back or they may expect some reasonable percentage in return. Now, whatever helper C did to B is called as maintenance and champerty. Now, why is this opposed to public policy? It is good only, no? Remember, maintenance and champerty, if they are reasonable, it is legal and it is not opposed to public policy. If maintenance and champerty becomes unreasonable, maintenance and champerty becomes opposed to public policy. If it is unreasonable, I give you money now. Give me 25% of what you win in the case. That becomes unreasonable. In such case, people maintenance and champerty becomes opposed to public policy. And when else it will become opposed to public policy? Now, my question, why is C helping B? Because C wants to take revenge against A. So I'm helping you not with a good intention. I'm helping you with a bad intention. So my intention is bad. In law, we call it as malicious motive. Malicious means people bad. So if the reason of a person helping you is bad and not good, we call it as what people again opposed to public policy. Understood this whole part? All of you? Clear? Yes, sir. Okay, the last part, sir. Wagering agreements. What do you mean wager, pa? Wager. What is wager? Wager. Betting. Yes, sir. Anything which is gamble is called as people wager. Are wagering agreements valid, invalid? What do you think? They are void. They are not enforceable in the court. What do you mean by that? Let us imagine I purchase a lottery ticket. I win. But if the other party does not give me money, I cannot go and fight this case in the court. Court will not help me to recover money. Same is the example for all the gambling related activities. If you win, if the other party does not give you money, you cannot enforce it in the court. Understood all of you? That is only called as what? Wager. Wager is nothing but people gamble. Agreed? So nothing but it depends upon an uncertain event. You can never predict it. You may win it, you may lose it. Such things are called as what people wager. Now, transactions which are similar to wager, lottery transactions. So, lottery transactions are illegal in India and hence it is even punishable. Now, in class, I would have said 100 times here. Remember, we are only seeing from Indian Contract Act point of view. But for this wager, that is lotteries, there are lottery comes under state specific. Remember, union is stateless. Lottery is a state list matter. That's why people, anyone from in Karnataka, do you see lottery tickets? Anyone from Kerala? Lottery tickets valid. Every shop you guys can find it. In fact, the government only runs the lottery in Kerala. It's a state specific matter, but we are only seeing it from Indian Contract Act point of view, and hence I'm telling you it is illegal. But not, this is not a, I'm saying for your marathon, this much is sufficient. Read and go illegal, that's all. But if you guys get confused and all, how sure in my state it is valid, if that is the case, then Goa working only on gambling, casinos, highest and biggest revenue for the state. You need to have a license to run it. Then how come the entire state is running? It's legal there. Agree? It's a state specific law. So there it is valid. Clear all of you? Hello? Okay. Lotteries are illegal in India and hence punishable. What if the lottery is run by government? It is still considered as illegal only. But the government cannot be punished for this. Example I told you, no? State of Kerala. They only run it. then we will not punish it, but still it is considered as wager only. It is void. Clear? Yes, sir. What if it is a crossword puzzle? If it's a crossword puzzle, now what is crossword puzzle? Your Sudoku, whatever. Now my question is, how are you deciding the winner? Is it depending upon the skill or the luck? What do you mean by that? Imagine I will conduct one crossword puzzle inside the class. I'll keep one box here, put all your solutions here. I will shake it. I'll take one. Whoever wins it, now they will get the prize. Did you win because of your skill or luck? If it is luck, people, remember it will be considered as a wager and hence it is void. Sir, no, sir. I will say, people, I'll give you 10 minutes. Whoever comes and presents your answer first, they will get the prize. No, a person won it because he was fast. And you won it because of your skill. Now, second question. Okay, you won it because of your skill. What is the cash prize? If the cash prize, people, if it does not exceed 1,000, up to 1,000 rupees and skill, then the contract is valid. Sir, if it is based on skill, but if the cash price is 2,000 rupees, then you will treat it as void. Is clear? Yes, sir. Next one, speculative transactions. What are speculative transactions, people? Nothing but you can imagine share market transaction. If you are doing it inside the system, like as per the law, open a demat account, trade it normally, that is considered as valid legal transaction. Now, for example, you guys do not have a demat account. Now, what will you guys do? Outside the system, you guys are settling. Meaning, I'll say, Macha, better. Share price of Infosys is 1,500 today. By this month end, the share price will go to 1,750. It's a bet. Where are you doing it? Not inside the market. You're doing it out of the market. This is considered as what? Wager. Inside you do it, it is valid. Outside you do it, it's a wager. You cannot do it privately amongst you. Do it inside the system. Clear? That is called speculative transaction. Next one is people horse race. What is horse race? Horse race, people, is nothing but you have your jockey and all that is all. That is called as what, people? Horse race transactions. If in a horse race transaction, people, if the prize money is less than 500, it will be considered as wager. If it is more than 500 people, it is considered as valid. Generally not required. The logic here is, people, a person who is betting less than 500, you do not know anything about that particular game. A person who is betting more than 500 is knowing something about the game. Like, I know how the horse is built. I know the past performance of this rider. I know everything. Only then I will invest more than 500. And I'm telling you, in 1872, it is 500. Yeah. In 1971, my father's salary was 500. 100 years after that, I'm telling you. You can now what is the value of 500. Yeah. So it's a huge amount. In 1872, 500 is a huge amount. Yes. So less than 500 was considered as wager, more than 500 was considered as valid because it's a conscious decision. So I'm saying a lot of money if you're putting, that means you are a person who is literally in control of that game. You're not coming it like an outsider, like we do know CSK versus RCB. Yeah, I'm talking from the owners of CSK versus RCB now. Imagine they are coming. That is valid, not us. That's what is the scenario here. Clear? Huh? Understood? Huh? Okay. Transactions resembling wager but are not void. Chit fund, something similar to wager but not void. Not required for us. What is chit fund and all? They'll not ask you. Share market transaction, I told you. Inside the system valid, outside the system void. Game of skill, crossword puzzle, provided the prize money does not exceed 1,000 rupees. Contract of insurance, when we are doing indemnity contract, I'll tell you what is this. Is clear all of you? Okay, chalo, today we'll wind up. For tomorrow, we might take a little more. Yeah, be prepared and come. Clear? Tomorrow we'll do some more questions also. We'll take more questions. Let us quickly see some questions that we did yesterday. That is, we had done some units. So let us do the questions first and then let's start the class. Dana. Okay, start. Explain the type of contracts in the following agreements under the Indian Contract Act 1872. A coolie uniform picks up the luggage. A coolie in uniform picks up the luggage of A to be carried out of the railway station without being asked by A, and A allows him to do so. What type of contract? Implied contract. Obligation of the finder of lost goods to return them to the true owner. What type of contract? Quasi contract, huh? Yes, sir. Quasi contracts. A contract with B, owner of the factory, for the supply of 10 tons of sugar, but before the supply was affected, the fire caught in the factory and everything was destroyed. What type of contract? Void contract. Very good. Okay, next one. State with reasons whether the following agreements are valid or void. A clause in a contract provided that no action should be brought upon in case of breach. What type of can we have this clause? A clause in a contract provided that no action should be brought upon in case of breach. What is the provision?
They should not contain any
Opposed to public policy, but what is the main heading? What does it come under?
legal procedure.
Agreement in restraint of legal proceedings. No one can stop you. Now, for example, imagine in invoice of ArivuPro, we clearly put a point. If Arivu does not do a class because of any reason, you cannot go to court. Can we add such points in your agreement? Even if it is added, it will be considered as void. No one can take away your legal right to go to the court. It is your right. Even if such agreements are there, even if such clauses, clause means what? A paragraph. Even if it is there, it will be considered as void. It's a void agreement. Here, no one can take away your legal right to go to the court. It is your right. No one can take it away. Even if you have signed it, no one can take it away. That's the point. That's a provision. Clear? Restraint of legal proceedings. That cannot happen. Okay, next one. Where two courts have jurisdiction to try a suit, an agreement between the parties that suit should be filed in one of those courts alone and not in the other court. Is it a valid agreement? Void agreement? So let us imagine in Bangalore there are two courts. There is an agreement that we should take this court, whatever the case between us, we should be taking it only in court A, not in court B. Such agreement between the parties, is it valid, void? What do you think? Hello, good morning. Void, voidable. Valid, void, what do you think? I hope you guys are understanding the question. There's a dispute between Arivu and you. Now in Bangalore, there are two courts. We are saying that if there is any dispute, we need to go to the court in Jainagar, which is nearby. And you guys have also signed this agreement. What will happen to such agreements? Is it valid, void? What do you think? Valid? It's a valid agreement. It's not stopping your right. No. Just that between two courts, you're choosing one court. It's a valid agreement. It's not void. It's a valid contract. Agreed on? Next one. X offers to sell his Maruti car to Y. Y believes that X has only a Wagoner car, but agrees to buy it. What type of agreement? Void. Void agreement. Valid agreement. Read once. Huh? Voidable. Void ab initio. Under what grounds? Consensus ad item. Also, it can be mistake of fact, bilateral mistake. Both of them are under a mistake. That's why it's a void agreement. What if it's a unilateral? That is only one person is under a mistake. Then it will be valid agreement. Yesterday we saw mistake of fact. You remember? Mistake of fact can also be considered as consensus ad item. It can also be considered as offer is vague and not certain. This answer can be written as those 3 points also. Understood? Okay, next one. X, a physician and surgeon, employs Y as an assistant on a salary of 75,000 rupees per month for a term of 2 years. And Y agrees not to practice as a surgeon and physician during these 2 years. Valid? Can someone stop you from doing business? Is it possible? Possible, lah. So, agreement in restraint of trade, you have to write those points. It is a reasonable restriction, hence it is valid. I'm only stopping you for 2 years. It's valid. If someone is stopping you forever, then it becomes void. Hello? Pakka na? Okay. Next, we have seen this, huh? Mr. B makes a proposal to Mr. S by post to sell his house for 10 lakhs and posts the letter on 10th April 2020. And the letter reaches Mr. S on 12th April 2020. He reads the letter on 13th April 2020. When is the offer complete? 13th. Whenever you get to know the knowledge of it, not when you receive it. Mr. S sends his letter of acceptance on 16th April 2020. Letter is put in post upon 16th April. And the letter reaches B on 20th April. On 17th April, S changed his mind and sent a telegram withdrawing his acceptance. Telegram reaches Mr. B on 19th April 2020. Examine with reference to the Indian Contract Act, on which day the offer made by Mr. B is complete. 13th April, that is whenever you read it. Okay, fair enough. Next one. Discuss the validity of acceptance. Is validity of acceptance. Is it valid, invalid? What happens? Can I withdraw the acceptance? Is it possible? Possible? Because people, when is the acceptance complete? From the acceptor's point of view, whenever the proposer reads it, here when will he read it? On 20th. When is he withdrawing his acceptance? 19th. So whichever reaches first, it will be valid. So 19th it is reaching, withdrawing. So acceptance, withdrawing of acceptance is valid. Agreed? Yes, sir. Okay, next one. What would be the validity of acceptance if letter of revocation and letter of acceptance were received together? Acceptance and withdrawing, both are reached on the same day. What happened? Whichever he reads first will be valid. Again, you need to prove. I can say I have cheated also. I read this first. That is okay. But evidence prevails. Okay, yeah. Which one? They have asked 3 questions now.
Last question.
I'll show you've seen. Okay. Mr. Ramlal Birla was a big businessman of the city of Pune, having 2 sons and 1 married daughter. He decided to gift his one house to his daughter. For this purpose, he called his lawyers at his house and made a written document for such a gift. The lawyer advised him to get the transfer document properly registered. When they were both going for the registration of documents, they met with an accident and both of them died. Later, his daughter found the document and claimed the house on the basis of the document. Explain whether she can get the house as a gift under the Indian Contract Act 1872. Why? Okay, so whenever you're writing exceptions to quid pro quo, whenever the parties stand in a near relationship or based upon natural love and affection, a contract can be valid provided the parties stand in a near relationship and the document has to be in writing and it must be mandatorily registered. In the given case, as the document is not registered, she is not the owner yet. The contract is not yet complete. My conclusion will be whether can she get the house? Answer is no, she cannot get the house. Here the word gift is misleading. Whenever the parties are in a near relationship, that too if it is a property, it cannot be on a oral basis. It has to be writing, it should be registered. Getting the point? Because in exceptions to quid pro quo, you have gift option also. There, all these conditions are not there. There are high chances students will write it as per that. Always remember, where will you get confused? The question will always have hints. Yesterday also you had a doubt between one question. Sir, why not that? Why is it this? The question will always have hint. That is, now for example, let us imagine this question, you are confused between gift and natural love and affection. Which one should I choose? For a reason they are telling father and daughter. Point number one. For a reason they're telling you the document was written and not yet registered. Point number two. When you have so many hints, it is your duty to choose the provision which has all these words and not gift. Understood? Huh? So based on those grounds, I'm telling you, it is not gift. It comes under natural love and affection. Hello? Brains are working, kada? Working, sir. You madi it work. It'll take time. Winter, no. Okay. Mr. Sham, aged 58 years, was employed in a government department. Okay. Mr. Sham, aged 58 years, was employed in a government department. He was going to retire after 2 years. Mr. Dev made a proposal to Mr. Sham to apply for voluntary retirement from his post so that Mr. Dev can be appointed in his place. Mr. Dev offered a sum of 10 lakhs as consideration to Mr. Sham to induce him to retire. Mr. Sham refused at first instance, but when he evaluated the amount offered as consideration, which was just double of his cumulative remuneration to be received during the tenure of 2 years of employment, he agreed to receive the consideration and accepted the above agreement to receive money to retire from his office. Whether the above agreement is valid. Explain with reference to the provision of Indian Contract Act 1872. Huh? Valid? Invalid? Why? Tell me the provision. Hey, remember in Indian Contract Act, Sale of Goods Act, answer is simple, yes or no. And there are high chances you getting it right because it will be evident. You can clearly tell is a yes or a no. And remember, people, you will never get a mark for a right conclusion, but a wrong provision. Meaning, operation successful, patient died. Ian, what's the use? So you just write yes or a no. Even you know, I know. It's a fluke. They between two words, there are high chances you can get a right one. There will be never a mark given if the conclusion is right, but the provision is wrong. So even if your conclusion is right, yes, you wrote it correct, but provision is something else. A patient came to you for a kidney problem. You did a open heart surgery. How is it right? You did operation, correct only. For that, should I pay fees? So provision is wrong. The conclusion is definitely wrong. You reach the conclusion through a wrong operation. So definitely you will not get a mark. Not even 1 mark. By mistake also I will not give you. Yes, sir. Okay, na. Tell me, what is the provision? Trafficking of public offices, legality of object and consideration, lawful object, lawful consideration. Under that it comes agreements opposed to public policy. Under that it comes trafficking of public offices and titles. Someone got no. Okay, understood. Until that extent, if you are able to write, macha, no, valuator Kamal will argue. Yes, he will be impressed. Until that extent, you should be able to write your provision. Provision is right, macha. Half life settled. Yes, sir. That's the problem. Okay. Explain the concept of misrepresentation in matters of contract. Sohan induced Suraj to buy his motorcycle, saying that it was in a very good condition. After taking the motorcycle, Suraj complained that there were many defects in the motorcycle. Sohan proposed to get it repaired and promised to pay 40% cost of the repairs. After a few days, the motorcycle did not work at all. Now Suraj wants to resign. What do you mean by resign? Cancel the contract. Decide giving reasons whether Suraj can cancel the contract. Now, see the question once. Tell me. Why? Provision.
Sir, what is misrepresentation is not done. Yes, sir. Because the person slower mentioned that he knows that the motorcycle is damaged or in a state that it won't work.
Okay.
And second thing,
So according to this is not misrepresentation, is what you're saying. Okay.
the rule of carrying the acceptance.
Let the buyer be aware. Okay.
And we can.
So under those grounds, Suraj cannot cancel the contract. Okay. Any other answer?
We accepted the 40% of the difference. Acknowledge that.
But what, under what provision you are writing? Provision is estoppel. Okay. Huh.
It is a voidable contract, but he's already ratified it. Like he got the 40%
Provision misrepresentation only. Huh.
He already accepted for the 40%. Now he cannot cancel.
Okay. Any other answers?
He should accept the offer. Like he got the compensation,
Hmm.
so he can't cancel.
Remember, people, in this is the first word itself is misrepresentation. Question is misrepresentation. Then why did they use the word misrepresentation in the first place? Look at the question also. Explain the concept of misrepresentation. People remember one more thing in exams. Now, this was a 6 marks question. People have literally ignored this part. Where is this? This part. Literally ignored. They only wrote the answer for the second part of the question. The question will have 2 questions at times. Not every time they will give it to you. Spoon feeding will not happen every time. Now, I'm telling you, at least 40% of the people did not write the answer for what is misrepresentation. Definition was also asked there. First thing, second thing. Now, what am I telling you? Sohan induced Suraj to buy motorcycles, saying that it was in a very good condition. After taking the motorcycle, Suraj complained that there were many defects in the motorcycle. Sohan proposed to get it repaired. Now, see, here there can be 2 issues. One, was Suraj aware of, was Sohan aware of these mistakes, or Sohan was not aware of those mistakes? We have to take a call. Now, if he was aware of the mistakes, you can call it as a fraud. If he was not aware of the mistakes, you call it as misrepresentation. You guys will have that question. Now, you tell me, is the question having a hint? What is the hint? They are telling you it is coming up with misrepresentation. They are coupling it with misrepresentation. So I will write with an assumption that Sohan is not aware of the defects that were there in the bike. Agreed? Hello? Okay. Second one. What are they telling you? There were many defects. Many defects in the motorcycle. Now the question is, were there these defects? Were they identifiable, non-identifiable? Have they given in the question? If it is non-identifiable, then, or if the question is silent, you do not assume that these were evident mistakes. Don't assume. If it was evident mistakes, they would have given it to you in the question. Then caveat emptor will apply. Yesterday I told you there is a crack, laminate is put. How will you identify it? If at all it is identifiable, they will give it to you in the question. Do not assume that it was an identity. How can you assume that it is an identifiable defect? They have not given. Hello? So you will be writing it as it was. Why I'll tell you, why did I assume it is not identifiable mistake? Because when he went back, Sohan agreed that I will take care of those defects and I'll also bear 40% of the cost. If it was not, then why will he bear it? Even he was not aware of it. That's why he has agreed to, pay for it. Agreed? Now, people, in misrepresentation, there will be a point. What is that point? In a misrepresentation, once you have identified a mistake, now you have 2 rights. Option number 1, what? It's a voidable contract. Go and give back the goods and get back your money. It's voidable. Option 2, if at all you go and say that there are defects, if the party says, I will take care of those defects, I'll pay for it, and you agreed. Now, in this case, he agreed. 40% cost was taken. The defects was rectified. After a few days, again few more defects come. Now the party does not have any right over it. Voidable contract only will be at once. It is not forever. Now, first time I went back. There were defects. 40% he paid. Done. Your right of rescinding the contract ended there when you took compensation. So whenever it's a voidable contract, you will have two rights. One, I can return the product, get back the money. Voidable. Option two, when the other party is saying that I'll fix it, then you take it, but you will lose a right to cancel it in the future. You cannot cancel it again in the future. Where is all this written? It is written in misrepresentation only. Hello. Exam question, no? 6 marks, sir. Good, no? Okay, we'll see this. Total we did it, huh? Huh? We didn't do this. Okay. Mr. Saman, AC is not working, huh? Are we feeling cold, hot? Yen kata hai? Cold, ah? Little, at least let us tell them to put it in fan mode. If not AC. When you guys come to see the class and all, you will be impressed by seeing AC. But मैं AC बैठा था. You'll note, there are 5 tube lights. You imagine it. I feel like you're sitting in. Priyanka, ಸ್ವಲ್ಪ AC on ಮಾಡ್ತೀರಾ? ಸ್ವಲ್ಪ temperature ಒಂದು ಸ್ವಲ್ಪ 18 okay, 20? ಒಂದು 24 ಇಟ್ಬಿಡಿ ಪ್ರಿಯಾಂಕಾ. Outside only it's 18. Okay. Mr. Samant owned a motor car. He approached Mr. Chotu and offered to sell his motor car for 3 lakh. Mr. Samant told Mr. Chotu that the motor car is running at the rate of 30 km per liter of petrol. Both the fuel meter and the speed meter of the car were working perfectly. Mr. Chotu agreed with the proposal of Mr. Samant and took delivery of the car by paying 3 lakh to Mr. Samant. After 10 days, Mr. Chotu came back with the car and stated that the claim made by Mr. Samant regarding fuel efficiency was not correct and therefore there was a case of misrepresentation. Referring to the provisions of Indian Contract Act, decide and write whether Mr. Chotu can resign the contract in the above case. Misrepresentation. Can I do it or not? Is it a fraud? Is it a misrepresentation? What is the scenario?
They already said that the fuel meter and speed meter are working correctly, so he cannot receive them.
Under what provision? KV tempter. Okay. Any other provision? They machas, all of you. Okay, read once and answer. No, all fine, all good. Provision. Don't tell me conclusion. Give me provision. You have to first diagnose the problem. Any answers? Provisions? Mistake of fact. Okay. Mistake of fact. Okay. Misrepresentation. Okay. So voidable. Okay.
So you told the fuel meter and speed meter is working perfectly. Yeah, it may be.
Give me fraud. Okay. Yes, any other answer? Misrepresentation. Can I cancel the contract? So do I have a right? Can Chotu resign the contract? Yes? All of you? No? Yadana on there, no. He cannot cancel. Why? Which process, sir? Simple, sir. You don't know what, sir. In real life, this is how we'll do.
had done something to the car, maybe it was his fault.
Yes, sir. Now, what happened? Correct, correct. That is what. Now I'll tell you what is the scenario. No, no. See, that is okay. I'll tell you. That is okay. See, now in your previous case, for the defects, did they give you any hint there? I told you there will be a hint given. Now, what is the hint here? For a reason they're telling you, this person is telling that the car will give 30 kilometers per liter, is what they're telling you is the mileage of the car. With that, they're telling you that the car's fuel meter and the speedometer and all that parts are working perfectly and properly. So, what do you mean by that? It was a duty of the buyer to check before he buys. That's why they're telling you there was no defects there. Even if you have driven for some day, 3 lakhs are investing, you'll not drive, Ada. You'll of course drive. You will do inspection. So this is where I tell you, they will give you the hint. It will be there in the question. Now in the previous part, they said damages was there. Anything like this was given? No. When nothing is given, then don't presume. When they give you this is what is called hints. This is what I tell you. There will be hints in the question. It's a matter of misrepresentation, agreed, or of fraud. Let us imagine they have not said whether he did it intentionally or unintentionally, but towards them they are telling you misrepresentation. There was a case of misrepresentation. They have said, okay, let us assume misrepresentation only. But do I have a right to cancel the contract? Answer is no. Why? Because if I have acted diligently with ordinary due care, if I had checked, I would have got to know about it. I did not check. So on this grounds, I cannot claim misrepresentation. So I cannot cancel the contract. Question will definitely have hints. You have to get that. Hello? If you guys are feeling these are little difficult, remember I've taken those questions only. That's why I call this as tricky questions. I'm done with your regular questions in the class. That and all is done. I hope you're getting the difference. Don't think, sir, anything we are not getting. Hey, the questions are taken like that only. I'm not taken 5 formal questions and 1 difficult question. If there are 40 questions in this booklet, all 40 are like this only. Hello? Pakka na? Okay. We'll do this one question and go for the next part. Huh? Okay. Next one. Okay. Srishti, a minor falsely representing her age, enter. Okay. What is the answer? Answer is that only. I told you no. K-bait enter. He has to check. That's the answer. It's not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. Meaning, even if you have checked a little, you would have got to know about it. In that case, it is not voidable. Clear? Huh? Hello. Macha, here car can be replaced with, imagine a person wants to go and buy. Of course, long back they used to give such questions. They wanted to buy a horse, a pig, but the horse was affected with fever. Things like that and all they will give. Yes, sir. So nowadays very rarely they give. It will be almost on automobiles only because more relatable. Agreed, but the question and answer is same. Okay. Anyways, see, Srishti, a minor, falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Gupta, owner of SP laptops, for purchase of laptop on credit amounting to 60,000 for purchasing a laptop on 1st August 2021. She promised to pay back the outstanding amount with interest at 16%. 16% per annum. By 31st July 2022, she told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay it back on her behalf. After 1 year, When Srishti was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she was a minor and now he couldn't recover a single penny from her. She will be an adult on 1st Jan 2024. Only after that agreement can be ratified. Explain in which of the following ways Mr. Gupta will succeed in recovering the outstanding amount with reference to the Indian Contract Act 1872.
No way.
Huh. Huh.
Cannot, minor can say that there is a minor.
Minor can plead minority.
Then it cannot find this,
Correct. Minor can never bind parents or guardians. Minor?
cannot be, non-negotiable.
Okay. Minor agreements can never be ratified. Okay.
Cannot be as that for the money.
And yes, the main provision is minor agreements are void ab initio. So on all these grounds, I cannot recover the money from this person at all. Agreed? Yes, sir. Hello. Okay.
They're also in case required money from only for his base.
Necessaries. Correct. If it is for necessaries, yes.
Why do you think that? Or provide a markup for education?
Yes, it becomes necessary. So I think during COVID or somewhere they had asked that question because it was online education, right? They had used the word tab. There was a credit agreement entered with the minor for educational purposes, and the purchase was a tab. So is it recoverable? Answer is yes. It's a necessary now.
But from the property of the minor.
Minor. It will be from the assets of the minor. Minor will never be personally liable. So if minor has some property worth that much, that is tab only is there. No, I can recover that. Yes, possible. From assets. Clear?
She is falsely representing her age. Does it come under?
No. Because it comes under breach of contract only, this whole topic. Tort comes under, if at all your tort is a little different. So tort is clear. Tort topic does not include anything with regards to contracts. Anything other than contracts will be covered under torts. Yes, sir. Yes.
It is for the necessary. Then whether this guidance, the guardians provided or
No. Guardians are never liable, no matter what the scenario is. Minor will be liable, provided the minor has assets, even for necessaries. Yes. Here they can go on adding the question, what if there is a dependent on the minor? All that can come. Yesterday we saw the scenario also. For that also minor will be liable, provided they have assets. If not, no. Then the word you guys use is also called as minor's estate will be liable. Never write minor will be liable for necessaries. It's wrong. You have to write minor's estate is liable, because if estate is not there, minor will not be liable. So that is how important using the words will be. Clear? Hello? Okay. Let us go back to some chapter. Unit 3 was done, Noda? Okay. So take class till 4. Randomly, okay. People, unit 4 down. Performance of contractor. See, we'll take today one more thing on YouTube, that ArivuPro channel. I think past 5 or 7 RTPs, 7 MTPs. I've solved and I've put it on YouTube. There is a tutorial I've done and put it how to write your answer. And how I did not tell it orally. I have also written one answer, one whole answer. If there are 2 questions involved, how to write. If there is 1 question involved, how to write. That is also put. When materials are available and you do not utilize it, don't blame me. last attempt, I have put what are the important topics for the exam. Around 65 marks has come, and still we failed. Sir, excuses, sir. Only excuses, sir. And I think I had given what? Last time I think I had given the chart book also. Till date, one day I had not given. Full chart book I had given free of cost. This chart book on that Arivu thing only. Go and check that YouTube that link is there. Last time marathon link is there. Yeah. Whatever can be done from my end, I have done. Section lists or sections are difficult, sir. You don't know. I put everything under one and I gave provision. Every chapter wise, I have given section list. What else you want? Spoon feeding to maximum. Correct, Noda? Then I think 14 RTPs, MTPs put together is solved 2.5 hours. Just to play it, more than 150 questions right in front of you, more than sufficient for law. Because the questions will repeat, what more can they invent? For invention also there will be one dead end, no? Yes or no? So make use of all of that. Okay. One more thing I've not, last time I did one more thing also. The entire case law compilation, your entire CA foundation laws, even if one letter case law is there, I've recorded and put it. 2.5 hours video. More than, I think, around 100 cases has been discussed and put it on YouTube. Put case laws, CA foundation law, you will get that video. And still we complain. Yes or no? ಏನಿಲ್ಲ ಅಟೆಂಪ್ಟ್ ತೋ ಝೀರೋ ಏನೋ ಎಫರ್ಟ್ ಇರಲ್ಲ. You're getting how much the what more you want. I am not writing your exam. That's the only thing pending. Okay, see here. In this year, this is 4th marathon I'm doing for CA Foundation. In law, nothing will change. That marathon only can run. Sir, we want marathon, sir. Noda? Okay. Notary. Performance of contractor. There are two types of performance exams. One is called as actual performance. One is called as attempted performance. Now, what do you mean by actual performance? Actual performance is nothing but where the obligation of the parties come to an end. Nothing but executed contract. I said I will teach you. You said you will pay. Done. Everything is done. It's called as actual performance. What do you mean by attempted performance? When one party makes an attempt to perform, but the other party is not willing to accept it, it's called as attempted performance. Example, Flipkart makes an attempt to deliver. You are here. Who will deliver? I mean, who will receive it? If someone is there, yes, they would have received it. What if no one is there? You will get a message. Flipkart has attempted to deliver. That is only called as attempted performance. Hello. Continuing, I'm just connecting one more topic here. Sale of Goods Act. Whenever basically a seller has attempted to deliver, and if a buyer has not received it, now the seller will take back the goods. The seller has it. If any damage happens to those goods, that will be at the risk of the buyer and not at the risk of the seller. Connecting those two topics, just telling you. Yes? What is the effect? The promisor is free from any liability. The effect of refusal to perform, the other party may put an end to the contract. Flipkart can say, go to hell. I will not deliver. They have a right. I will deliver. I'll try to deliver once. If you are not accepting it, I have a right to put an end to the contract. But always, I'll always tell you the first point I tell in the classes, Indian contract, sale of goods act, partnership are all private contracts. You guys can have your own clauses. When you guys have not agreed anything is when these contracts will apply. So in Flipkart, they have clearly agreed. We will Sir, we will come second time, third time we will come. They are okay. But what if there is nothing agreed between you guys? That is when Indian Contract Act will apply. Understood? Hello. Okay. Who can perform the contractor? First one, who can perform the promiser himself? When can promiser himself perform? Whenever the contract says so. I want you only to perform. I don't want anyone else to perform. When will this scenario come into picture? Whenever there is any skill, confidence, talent involved. It can be an artist, it can be a singer, it can be an actor. We want you only, sir. We don't want anyone else. If that is the case of the contract, who can perform? Always the party himself has to perform, no one else on his behalf. Agreed? Sir, what if that is not the case? What if there is no personal skill or confidence involved? Then anyone else on his behalf can perform. Hello? Sir, that is what? Let us imagine A has taken loan from B, 1 lakh. To repay loan, you want special skill and talent. No, A dies. Now, who will have to repay the loan? It has to be the legal representative. C will be liable to pay the money to B. Sir, A agreed to sell one, what do you say, art, a picture, a canvas painting. I agreed to draw and I agreed to sell, and A died. Now C is liable to draw it again. I will draw, but I'm not sure whether it will be your picture or not. Now, am I liable? Answer is no, because there is skill and talent involved. So I cannot hold the legal representative liable. In such case, what will be the effect of the contract? Whatever advance I've taken, I need to give it back, and the contract becomes void. It's a void contract. Agreed? Supervening impossibility, death of a person. Okay. Legal representative, whatever I told you. Personal skill involved, legal representative not liable. If it is personal skill not involved, legal representative is liable, provided up to what extent? A has taken 1 lakh rupees loan. A passes away. C is liable to repay. C is liable. To what extent? So C has got some inheritance. Assets I would have got, no. Whatever is the value of the assets I got, only to that extent I'll be liable. If I got 50,000, I'll be liable for 50,000. I got 5 lakh. Then I'll be liable to pay this 1 lakh. Agreed? Okay. Next one, people. Agent. Of course, we'll be seeing in the agency chapter. I can appoint someone else to act on my behalf. Example, real estate, car. In all these cases, you are not going and selling and buying. No, you have a mediator. They are called your agents, representatives. Allowed. Possible. Next one is third person. Who is the third person? Someone acting on your behalf is called as what? The third person. Generally, who will this be? Brokers. Now, whenever a person is specifically appointed, we call that person as an agent. Whenever a person is not specifically appointed, we call such person as a third person. Now, how do we say that, sir? Now, for example, old lady, brother, there was a daughter. Now, old lady gave the property, but the contract was between these two people. Agreed? Now, the brother did not appoint the old lady to do anything, but the old lady gave the property. On that basis, the brother is entitled to get a pension from that KD. Agreed? Now, there you saw this rule. Consideration may move from promisee or any other person. Any other person is a third person. Now, I did not appoint her. Did I appoint her? No. She did it on her own will. So, third person is never appointed formally. Like an agent, those words will not be used. Hello? For example, people, there was a contract between A.R. Rahman and PVR that I will come and perform on a particular day. But A.R. Rahman could not come. A.R. Rahman sent Anirudh. And PVR was okay with it. For them, the life is still going on. Special skill and talent only. But I'm saying they had a right to cancel the contract. They could have said, no, we don't want Anirudh. But they accepted Anirudh. Now this is called as third person. Now they cannot cancel the contract in the future. Hello? Understanding? Yes, okay. Third person. If third person performs, he cannot afterwards enforce it against the promiser. Anirudh performed. Now you cannot go back and hold A.R. Rahman liable. When he came itself, you have a right. You can say, no, 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 sir, you only should have come. We will not accept Anirudh. You can stop. But once you accept it, you cannot again, you cannot again cancel the contract. You cannot again ask for compensation. All that not possible. Even when such act is not authorized by the promiser. So even if I have not appointed you, if the other party did it on their own, it will still be valid. Chinnaya versus Ramaya. Okay, last one is called joint promises. What do you mean by joint promises now? When two or more parties together agree to repay something or perform something is called as what? Joint promiser. A, B took a loan from C. How much did they take? 2 lakh rupees. A took 1 lakh, B took 1 lakh. Now when they have to repay 2 lakhs only. Now in this case, what will happen if A becomes insolvent? How much should we repay? If A becomes insolvent, together we have taken 2 lakh. Now A has become insolvent. How much should I repay? 2 lakh only. Who will repay? A's legal representative along with B will have to repay this 2 lakh to C. Because whenever there is a death, the next rule that will apply is legal representative. Legal representative will be liable to repay the money with the other joint promiser. Sir, what if A does not have legal representative? No assets, nothing. Then in such case, people, it will become B's liability to repay the entire 2 lakh. Agreed? That is what is the rule of joint promisers. Exam point of view, there can be a question. Remember and go. Clear? Understood? Any doubted? Whenever there is a contract of joint promise, what is joint promise? When two parties or more, let us imagine 3 parties are there. Together they borrowed 3 lakh from one person and each person has taken 1 lakh in that 3 lakh. Now if one person dies, now what will be the liability? Is that person exempted from repaying? They're telling you whenever a person dies, their legal representative will have to pay the 1 lakh along with the other promises. Sir, what if even legal representative is not there for this person? In such case, what to do? That the other 2 joint promisers has to share that equally. They may ask you a question in this way. How will they share the liability? It will be shared equally. So they'll be liable for 1.5 lakh each. Clear?
Like what if the legal head only now 50,000, the ability to pay 50,000?
Then, now, for example, if legal representative is there, if legal representative is able to pay 50K, then rest of the 50K will be paid by these 2 people. End of the day, they will have to pay 3 lakh and legal representative is liable to the extent of the assets they got. They will be liable. Clear? Okay. Same rule will apply. Let us imagine if B became insolvent, then the entire liability will now be on C. Now, how much will he pay? Let us imagine the legal representative of A has only 50K. See, your answer always ends whenever there is an insolvent. A solvent joint promiser will always have to bear the loss. How much ever it is, I need to pay. There your answer ends. But in reality, if you ask me, I cannot recover. But if I want to recover, the insolvent will have to file an application to the court saying that, sir, I am no longer insolvent. Please treat me as solvent. The court will remove the tag put on you. They will remove that insolvent tag, provided they have a condition. The condition is whatever liabilities you have to repay, first to repay. If you're able to repay, now the tag put on you called as insolvent will be removed. Yes, sir, but not required for your exam. Then, okay, this is joint promisers. What is joint promisee? When one party is taking something from more than 2-3 people, is called as what? Joint promisee. So I am promising for more than one party that I will repay the loan, not with one person, with more than one person. Then such type of loans are called as what? Joint promises. Yes, sir. Example, where can this happen? Vijay Mallya's case. This type of borrowing is called as what? Consortium lending. Consortium means what? We are giving money together. Vijay Mallya borrowed money from how many banks? SBI was the lead bank. Lead bank, meaning application came to them. From them, the application went to another 4 or 5 banks. Punjab National Bank, Axis, ICICI, HDFC. There are many people involved. Together, they gave loan. In one application, that is important. Not many applications was not there. They were all part of one application. Such type of loans we call as what? Consortium lending. Not required for us. But all these banks put together, we call them as joint promises. Huh? Promisee. Promiser is a person who is promising. Promisee is a person to whom it is being promised. Clear? Hello? Okay, done. Next one, joint promises. Rules of joint promiser. What are the rules? Any one of joint promisers may be compelled to perform. Agreed? I can ask one joint promisers to repay the entire debt. Agreed? He can later recover from the other joint promisers. So let us imagine there was A, B, C. We have taken loan from D. D can compel only A to repay the loan. Yes, A will be liable, but A can later recover it from B and C. That is what is the next rule. Correct? Okay, next one. If any joint promisers makes default, remaining joint promisers will bear the loss. Your example, insolvent. Next one, even if one of the joint holder is released by promise, he continues to be liable to the other promisers. Meaning what? If there is A, B, C, and there is D. If D tells C, I will not recover any money from you. You go. I will recover the entire money from A and B. You have waived C from his liability. You have taken entire money from A and B. But A and B can recover the money from C. D might have exempted you, but you are liable to the other joint promisers. C is liable to A and B. Clear? Okay. If any of them dies, what will happen? The legal representative will be liable with the other promisers. Agreed? Okay, done. Joint promise we saw. Time and place of performance of the promise. Where will the promise be always performed? If time is not specified, if place is not specified. In such case, what do we do? It will always be performed within reasonable time. What is reasonable is always matter of fact. It depends upon product to product. Sir, where will we perform? The promiser should ask promisee where to deliver. If nothing is agreed in the agreement, then in such case, the promiser, Flipkart will ask, sir, where do you want me to deliver? If nothing is agreed. Sir, if time is specified, place is specified, then the promise will be performed at that time, at that place. Sir, if time is not specified, if a place is not specified, but the application is to be made, that means what? It is a buyer's responsibility to ask, sir, can you please deliver the product to me in this place at this time? It is my responsibility. Agreed? Yes or no? See this if you guys have any doubts. Let me know. What is this place and the time of performance? Now, for example, you guys go and buy one grocery items in a nearby shop. You buy something nearby shop. You tell me when should that shop person give you the grocery items? And at one is time, one is where, and one is when. Tell me, first scenario, where will the shop person give it to you? He will give it to you wherever you have entered into a contract. But let us imagine people, the shop person agreed to deliver. Sir, you go home, sir, we will deliver. You tell me, where should I deliver? What time should I deliver? Now, that is what we are seeing. If between us, we have agreed where to deliver and what time to deliver. If we have agreed, it is a duty of the shopkeeper to deliver at that time, at that place. Sir, what if nothing is agreed? What if nothing is agreed? That is what is given here, not specified. Time is not specified, place is not specified. In such case, what will we do? Now, it is the responsibility of the shopkeeper, promiser, to ask promisee, sir, where can I deliver? Where do you want me to deliver? Tell me, sir. Now, people, by default, where will I give the goods? I'll give it in the shop. Agreed? Hello? Sir, no, sir. I have clearly written the home delivery is available, but you need to ask for it. Home delivery is available. By default, I will give it in the shop only. If you ask for it, I will deliver. It is written in the shop. Now it is whose responsibility to ask the shopkeeper to deliver? It is a buyer's responsibility. That is what is this. Application is to be made. I need to ask for it. If time and place, nothing is agreed. By default, I will give it in the shop only. But if it is clearly written on the top, upon request, the home delivery is available. It is a duty of the buyer to ask for it. That is what is given here. Promisee's responsibility to make an application. Make an application means what? Ask. Understood? Hello? Okay. Next one. Next topic is called reciprocal promise. What do you mean by reciprocal promise? Yesterday only we saw. What is reciprocal promise? If you will do, I will also do in the future. People, what is that? Reciprocal promise is nothing but people bilateral executory contract. A and B both are agreeing today. A is agreeing to deliver the product in the future. B is also agreeing to pay for the product in the future. But both of them are entering into an agreement today. We call such type of contracts as what? We call such type of contracts as executory bilateral contract, and also it is an example for reciprocal promises. Example, you enter into a contract with Amazon for cash on delivery. Amazon tells you, I will deliver the product on 1st of Jan 26. You will also say, I will pay it on 1st of Jan 26. But the contract is entered today. Now, such type of contracts are called as what? Reciprocal promises. As on today, we entered into a contract today, no? But obligations of both the parties are pending. That's why we call these contracts as what? Executory contract. How many parties obligation is pending? Two. That's why we call it as bilateral executory contract. This is where I told you bilateral executory contract and reciprocal promises are same. Hello? Clear? Okay, now they have given you some rules regarding reciprocal promise, children rules. Now what is that? Promiser not bound to perform unless reciprocal promisee is ready and willing to perform. The Amazon guy has come to your home to deliver your phone. He will not deliver your phone until you are ready to pay the money. Agreed? That is what is given here. Promiser is not bound to perform. Amazon guy is not bound to deliver unless the reciprocal promisee, that is the buyer, is ready and willing to perform, ready to pay. If you are not ready to pay, he will not really deliver. Children rule. When one fails to perform his promise, he cannot compel other party to perform. Agreed? Sir, Amazon has come and what is that? The B is not willing to pay. I'm not paying the money, but I'm asking A to deliver the product. Will it work? Answer is no. That is what is given here. When one fails to perform, I did not make the payment. He cannot compel. I cannot ask Amazon guy to perform and claim compensation. I cannot tell him to deliver if I'm not willing to make the payment. Hello? Children rule. Order of performance. Who should give the payment and who should give the product? Order of performance means what? Amazon guy has come. Who should first give? You should give money and he will give the goods, or he will give the goods and you will give the money. What is the contract? What is the order? They're telling you, go as per the contract. Generally, they will not give you the product. If it is cash on delivery, they will check. What if fake notes are there? They will first check everything until that the product will not be handed over to you. I'm not telling in children. I'm telling in, say, for example, if you have given, say, mobile, say if it's an electronic gadget, if you are giving cash, they will check everything. Only if everything is clear is when they will give you the product. So order of contract is clear. First you pay. If everything is good, then we will give you the mobile. Sir, what if nothing is agreed? Then you will go as per the nature of transaction. Nature of transaction means what, people? In that particular industry, there will be a pre-mindset. Follow that. For example, you go to hotel. If you're going for self-service, you first pay and then eat. If you go for service, you first eat and then pay. Correct? Huh? So it is all dependent upon the nature of transaction, which can differ from industry to industry if nothing is agreed. Simple? Hello? Reciprocal promises, which are legal in part, if they can be separated, legal part is always valid, illegal part is void. We saw yesterday the rice and weed. Liability of party preventing the event. Contract becomes voidable, entitled for compensation. What do you mean by this? The liability of party preventing the event?
Promising from
Can you give an example? Okay, liability of party preventing the contract becomes voidable, entitled for compensation. You're saying Flipkart guy comes to your home, you are at the home. Okay, attempted performance. Okay, makes sense. Huh? Any other example? Okay, fair enough. Yes, both are correct only. Let us imagine now this furniture here, this was made by an order. So what do? We give a carpenter, we tell him that we want, probably some 40 benches to be made. We have two ways to do it. How? I will call the carpenter to the premises. I will tell, you tell me how much of wood you want. I will order it from some other place. Your job is to just come and do the benches. The material is mine. Yeah. So now what is happening? There is a contract between me and the carpenter. The carpenter comes the next day. He's in the premises. But people, it was my responsibility to supply wood. I was not able to get the wood on time. He has come. I have not come. I have not come with the wood. Now, can he perform the contract? Answer is no. That is what is the meaning of liability of party preventing the event. Meaning what? I have only stopped the contract. Who stopped it? I clearly said I will give the wood. Papa, that other party has come to the place. I did not supply the wood. So I have only prevented the contract. Now, in this case, what right does the carpenter has? Can the carpenter just go back or does he have any right? They're telling you they have a right. What? He can say, I am done. I will cancel the contract because from tomorrow I have a different contract. I cannot come again tomorrow. Next one, people, I can also claim compensation. What is claim compensation? I've come today, whether I work or not. It is your mistake. You have to pay me the labor. That is what is this particular scenario. Understood? Huh? Hello? Pakka? Okay. Next one. The same example can come one more place also. Negligence. Same scenario will repeat. Okay, next one. Impossible act. What is impossible act? Anything which is agreed to do an impossible act, people. If it is initially impossible, you will always treat it as void. Later on, impossible. Void agreement, void contract. Initial impossibility, void agreement. Subsequent impossibility, void contract. Change of law, alien enemy, destruction of subject matter, death. All that becomes void contract. Next one is effect of failure to perform. If time is essential, if time is not essential. What is this? Time is essential, time is not essential. So you would have ordered a product. At times, you do not mind. If the product is delivered now, today, or tomorrow, you don't mind. But there are some contracts where the product should be delivered within that time. When will that happen? Now, say for example, you want to, in example, I mean, in class we would have seen what? Where is time is essential? Imagine you guys would have given an order. You want to stitch a particular cloth. Yeah. Imagine you want to get married. He said, ah, yeah, waiting, sir. Now, people, so you want to get married. Now, he has given an order for probably a suit. Yeah. Now, they said, sir, we will deliver you the suit within next 5 days. Now, you tell me, people, in this 5 days, if they do not deliver, they said, sir, because of some technical issue, we could not deliver. On that wedding day, Papa, he is waiting for the suit. Suit did not come. So whatever dress he had, that only he had to get married. Now, people, next day he came and said, we are so sorry, sir. Here it is, your suit. Now, tell me, will he take the suit or not? Why? What will happen? One day there is a delay. For that, you can't adjust. What, in that one day you would have become fat or what? No, it will still fit you. A contract where time is essential. The time here is wedding. You are bound to give the product on time. If you do not give it, then what is the right I have? I can cancel the contract. The suit can be 20,000. I will say I will not pay 1 rupee. And not only that, you have affected my mental status. Yeah, the state of mind, I'm going for a toss. You might go very well go for a depression. Now, in that case, you can also claim compensation. So remember, whenever time is essential, you can cancel the contract as well as claim compensation. Whereas when time is not essential, what do you mean by that? Whenever you guys are ordering your clothes on Amazon or Myntra, you're doing a casual shopping. Now, if I ask you the purpose, no purpose, casual shopping. Now, in that case, is time essential? Answer is no. You do not have a right to cancel the contract if it is not delivered within the set time. Meaning, he said the delivery will happen in 3 days, but it delivered on the 4th day. At times it happens, a lot of times it will happen. Now, if it is not making any difference in your life, is it essential or not is what we need to check. If it is not essential, time is not essential, then you do not have a right to cancel the contract, but you can claim compensation. So time is essential, time is not essential. If time is essential, you can cancel the contract, you can also claim compensation. If time is not essential, you cannot cancel the contract, but you can claim compensation. Clear? Hello? Okay. Next one, people. Appropriation of payment. What is appropriation of payment means? There can be a question here. Remember, important. What do you mean by appropriation of payment? Whenever a debtor has taken multiple debts from the same creditor, I've taken 1 lakh, I've taken 3 lakh, I've taken 35,000 on January, on March, on May. Now, when A is repaying the debt, when A is paying the debt back, when A is repaying the debt back to B, when A is repaying the debt back to B, now you tell me what is the order of payment. First, the debt was taken in Jan, one was in March, one was in May. The first option is always given to the debtor to choose which money you are repaying. I can choose whether it is towards the repayment of first loan, second loan, third loan. it is always at the option of the debtor first. Sir, what if debtor is silent? Now what will happen? Now the question is, how much did A repay? A repaid 35,000, but A did not specify towards which transaction he is repaying. Now you tell me, towards which transaction you will take? First, second, third. Third. This is only called as what? Circumstances. I am repaying 35,000, but I was silent. But exactly for 35,000, there is one more debt. Then the circumstances say that I am repaying the debt for the third transaction. That's the second scenario. First will always be people debtor. Second people is circumstance. Sir, now what if debtor is also silent? Circumstance is also silent. Now what to do? It is the creditor's choice. He can take it in any order. Sir, what if debtor silent, circumstance silent, creditor silent? Now what will you do? Always you will go in FIFO method, first in, first out. So you'll always go for the first transaction. Clear? Exam point of view, important. You can expect a question. Next one, contracts which need not be performed, meaning which are exempted. You can classify this into mutual agreement. What is mutual agreement? These contracts need not be performed, it seems. What do you mean by that? Meaning you have entered into a contract, later they're telling you, you need not have to perform this contract. What type of contract is that? First one is called as novation. What do you mean by novation? A and B had entered into a contract. For example, let us take this building only. We have entered into a rental agreement. Now, ArivuPro has taken this building on rent from this landlord. After 2 years, full vastu worked. We want to buy this location only. Now, people, we have entered into a lease for 5 years. But after 2 years, we feel that, this should not be rental anymore. The property is really working out for us. So what do? We decide to replace this by a purchase agreement. Now this type of contracts where we replace the terms completely, but we are doing it within us. We are replacing it. Now we call these as what? Novation. Novation means what? When one contract replaces by another contract. Such type of contracts are called as novation. For example, one more example. A came and did admissions with B. I mean, let us imagine. There is a person, student called as B. B came and took admissions with ArivuPro. But B, because of some reasons, B does not want to continue the course. But let us imagine if refund was not available. What will A say? Okay, you do one thing. In your place, you send any other student. That's okay. Now B will tell, okay, instead of me, I will send another person called C. Is it okay? Now we will say, okay. Now people, course is same, fees is same, the invoice is same, everything is same. But in B's name, we write now C. In attendance register, we'll write C. Now these type of contracts again is called as what? Novation. Why? In the same contract, only the party's name is changing. Everything else is same. You call it as novation. Remember, whenever the party's name change, it will always be called as novation only. Is this clear? Hello? Pakka. Sir, there is a contract between A and B. The loan is 1 lakh. Repayment is 2 years. Rate of interest is 15%. Now let us imagine this 2 years, we are making it 3 years. This 15%, we are making it 20%. Now what type of mutual agreement is this? This will come under alteration, change of terms in the existing contract. But name is not changing. The rest of the terms are changing. You call it as what? Alteration. Hello?
Yes, sir.
So going forward, the loan, it will no longer be for 15%. That is exempted. That need not be performed. It will now be performed for 20%. Agreed on? The third one is called as what? Rescission. What do you mean by rescission? Rescission means what, people? Cancellation. For example, the suit was not delivered on time. What will he do? When time is essential, he will resign the contract. If you give it to me tomorrow, I will not take it. The contract need not be performed. The contract will come to an end when time is essential. Agreed? Yes, sir. Okay. The last one is called as remission. What do you mean by remission? Remission means waiver, give up. Example, let us imagine Vijay Mallya had to repay to the banks somewhere around 9,000 crores. Vijay Mallya made a proposal. I cannot pay 9,000 crores. I will pay 5,000 crores. Can we settle this matter before going? I said I will pay 5,000 crores. I will settle this matter. Is it okay? If banks had agreed, you call this as what? Remission, waiver, settlement. Now going forward, let us imagine in the future, Vijay Mallya earns more money. He earned another 10,000 crores. Banks cannot go back and collect that rest of the 4,000 crore. You gave up your right. You settled once. That's all. That contract will come to an end. It will not be performed again in the future. So what are we seeing? When will a contract come to an end? When will the contract need not be performed? When the party has given up his right. I had a right to collect 9,000 crore, but I'm collecting 5,000 crore and I'm settling with it. I cannot demand the 4,000 crores in the future. That is called as what? Remission. Remission is also called as waiver. I'm giving up my right. I cannot collect the 4,000 crores in the future. Agreed? Understood? Okay. Last one, people. I told you, this is only called as promiser need not perform and promisee neglects performance. The carpenter example. Nothing but it is also called as negligence. Teacher gives everything. Student does not take anything. Negligence. Teacher is exempted from his liability. I am no longer liable for your result. I have done everything. Correct? No. Negligence is on the student's part. Hello. Again, carpenter example. Same thing will fit here also. Clear all of you? Hello? The last topics are discharge of a contractor. When will a contract will come to an end? First one, simplest one by performance. A delivered the product, B paid the money. The contract comes to an end. The parties are discharged. Next one is mutual agreement. Mutual agreement is nothing but novation, recession, alteration. Just now we saw. Next one is waiver, Vijay Mallya case. Negligence of performance, carpenter case. In these cases, contract will come to an end. The parties are discharged from obligations. Next one is impossibility by performance. What is this? Nothing but subsequent impossibility. Correct? That is the destruction of subject matter and as the case may be. Death. Next one, discharge by lapse of time. What is this lapse of time? I have to repay the debt within 3 years. If I don't repay, I have to go to the court within 3 years. If I don't go to the court within 3 years, court will not help me to recover the money. Legally, you are discharged. If he pays money, you take it, but you cannot go to the court and enforce the contract. Correct? Limitation. Time bar that we call no. Next one by operation of law. What is operation of law? Shoaib Akhtar. Change of law. Illegal, subsequent illegality. A person becomes alien enemy. India versus Pakistan. Government passes an order that going forward, do not enter into any contracts with Pakistan. What about the contracts already entered? That is only called operation of law. Parties are discharged. Shoaib Akhtar, of course, we agreed for 5 years. Within 2 years only, we took back. He can't file a case on us for compensation. It will be discharged. Contract will come to an end. Next one, breach of contract. Next topic we'll see. Next one is called merger of rights. What do you mean by merger of rights? That rent and thing I told. What is merger of rights? ArivuPro had taken a building on lease from B for 5 years. This is lease. After 2 years, Vastu worked. We wanted to buy the land. Sir, for 5 years there was lease. In the 3rd year, we are entering into sale deed, meaning we are buying the property. That means what? At current point of time, There is a lease agreement also, sale deed also. This type of thing is called as merger of rights. Now I am a tenant also as per lease agreement. As per sale deed, I am a owner. I am a tenant as well as owner. Merger of right means what? One person enjoys two capacities. It's called as what? Merger of rights. In that case, which agreement will prevail? Lease agreement or sale deed? Whichever agreement is superior will prevail. That is, sale deed will prevail. Lease agreement will come to an end. So this is what is discharged. Agreed? Hello? Pakana? Okay. Okay. Let's start the next unit. Unit 5, breach of contract and its remedies. Okay. We will see here breach of contract and its remedies. Now, what do you mean by breach of contract? Whenever there is a agreement, A agreed to deliver certain products to B. B agreed to pay some price whenever the products are delivered. Now, A is not in a position to deliver the products. He says, I'm unable to deliver the products. Now, what will be the effect of this contract? Now, this is only called as what? Breach of contract. Now, breach of contract can happen in two ways. One is called as actual breach, one is called as anticipatory breach. Actual breach is nothing but whenever the performance of the contract is happening during the performance. If a party resigns, he steps back. That is only called as what? Actual performance. For example, now let us imagine the class is going on. The class was supposed to be till 2 o'clock. The class is going on during the performance. I will say, people, let us discontinue the class now. Now, this is called as what? Actual performance. When the contract is happening, a party resigns the contract. That's called as what? Actual performance. So it will happen during the performance of the contract. The next one is called as people anticipatory breach. Tomorrow you have a class. I intimate today that people, let us call off the class. Now this is called as what? Anticipatory. I give you a notice in advance prior. That is only called as anticipatory breach. In both the cases, you will be entitled for compensation. But in anticipatory breach, there is something called what? What is the right you have? In anticipatory breach, let us imagine A has agreed to deliver some 1,000 shirts to B. Now, I have agreed to deliver this on 10th Jan 26. The contract was made on 1st Jan 26. Now, on 5th Jan 26, A is calling up B and telling that I will not be able to deliver the product because of whatever is the reason. I cannot deliver you the contract. So there is a breach of contract. I'm canceling the contract, whatever we have entered. Now I'm intimating it to you in advance, 5 days prior. Now, what is the right the B has? B has two rights. One, he can immediately cancel off the contract. Meaning, I will start looking for an alternative, because what if you give me the product in the future? I'll be bound to take it from you also, again from others also. To avoid that, what I can do, I can immediately cancel the contract. And what I will do, I will start searching for an alternative. Or I can give you some time. It's okay that trying. You have time till 10th, no, you try till then. Even on 10th, if you are not able to give, then I will cancel the contract. So you have two rights. One, immediately cancel. Next one, wait till 10th and cancel. Whether you immediately cancel or wait till 10th and cancel, you still have a right to get compensation. That right you always have, irrespective of the fact when you cancel. You still have a right to compensation. That is there. But always remember, the second thing will always come with one risk. What is that risk? So if at all on 5th Jan 26, he has intimated that I cannot perform the contract, I did not immediately cancel. I waited till 10th of January. Now let us imagine on 8th of January 2026, there is a fire breakout that happened in my factory. All my machinery is burst. Now, because of impossibility of performance, the contract will come to an end. It becomes a void contract, subsequent impossibility, destruction of subject matter. What is the difference then? Because the contract became void, you will lose a right to get compensation. That's the risk. because contract itself has become void. So the parties are discharged. Now you do not have any right of compensation. If you wait until the last day and if this happens. Of course, it is all one of a scenario, but I'm just telling you. I hope that part is clear. So you can either immediately cancel so that your compensation pakka you will get, or wait until the last day and cancel. So compensation depends upon if something happens, you will not get compensation. Clear? Understood? Hello? You guys are understanding it, huh? Okay. Okay, resigned immediately and claim compensation or wait and claim compensation. There is always risk of subsequent impossibility. And remember, people, impossibility is different from difficulty. What do you mean by that? Let us imagine on 8th of Jan, I agreed to supply of shirts. No, on 8th of Jan, let us imagine the cotton prices have gone up. I thought I can supply your contract within 1 lakh. But I did not know, I did not anticipate the raw material cost has gone up from 1 lakh to 1.5 lakh. Now, because of this reason, A is telling a subsequent impossibility. I will not be able to deliver the product on time because the prices have gone up. Now, can this be considered as void contract? Can this be considered as void contract? The cotton price, the raw material prices have gone up. No. Remember, this is difficulty of performance. It is your headache. You can't consider this as impossibility. There's a difference between difficulty and impossibility. I hope you're understanding. B will be entitled for compensation if you do not supply the product. Are you getting the point? Sir, now let us imagine A on 7th to 9th of Jan, A's workers went on a strike. Now, because of that, they could not manufacture the shirts. Now, because of that, he could not deliver it on 10th of Jan. Now, he's saying, hey, because of subsequent impossibility, the contract became void because my employees went on a strike. So, I'm not able to deliver the product. So, shall we cancel the contract? You will not be entitled for any compensation because subsequent impossibility. Can this be considered as subsequent impossibility? No, why? Because strikes or lockouts or nothing, whatever these things are, these are under your control. Remember, there is always a difference between impossibility and difficulty. These are all difficulties. Meaning, if, see, why will they go for a strike? Because they are not okay with some terms. Probably payment, they are not okay with it. They need an increase in pay. Now, if you increase the pay, they might have come back and they might work with you. Now that is called as difficulty. That's not impossibility. These questions can be asked in the exam. Impossibility is different. Difficulty is different. Strike, lockouts, commercially more. That is raw material prices going up. All these are difficulties and not impossibilities. And you cannot cancel the contract on that ground. You will have to pay compensation. Agreed? Understood? Okay. Yeah, I hope you all have already once at least studied Indian Contract Act. I mean, business laws. Huh? At least once. The marathon is becoming explanation. Da. Huh? You guys are not able to understand or I'm not getting it. The vibe is not there. Ah. Any of you, I mean, directly listening or reading it for the first time, complete law? No, all of you have studied at least once at least. Yes, you have a fair idea. Hello. Okay. Okay. Next one. Remedies. Remedies means what? What is the alternative I have? There's a breach of contract. Now, what do I get in return? A agreed to sell 1,000 shirts to B. Now, A did not sell it. Now, what is the remedy B has? What is the alternative B has? B has all these alternatives. What? First one is I can file a case for damages. Damages means compensation. Next one is rescission of contract. What do you mean by rescission? Resigned, meaning cancel. Because what if he comes and give it to me on 15th? So I do not want to take it because I'm looking for an alternative. So resigning of a contract puts an end to the contract. In the future, if you give also, I will not accept. I have that right. Next one, suit for specific performance. What is a suit for specific performance? When we are looking at minor agreements, I told you, I'll do this specific performance again. Now, what do you mean by specific performance? Generally, people, whenever a contract is entered, A agrees with B to sell one antique clock. Now, will I get this antique clock in some other place also? Answer is no. It's a rare model. It's a rare product. Now, if A does not sell this to B as per the contract, now B will file a case on A. I want the product. Now, he's not giving it. Now, if I go to court, technically, Contract Act means what? We saw yesterday, civil law, criminal law. Civil law, what is the remedy I am always seeking? What do I want? I need compensation. If money is given, my ego is satisfied. But remember, in antique items and all, money cannot satisfy your ego. That is one of a model. I want that only. Whenever a product has some specific importance, antique item, emotional attachment to you, those things cannot be compensated with money. In such cases, the court will order for something called as specific performance. So the court will say, no, 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 A, you can't give money to B. You have to give that clock only. That is only called as what? Suit for specific performance. I can demand for specific performance. In the shirts case, can B file suit for specific performance on A? Answer is no. The reason is, what special value these shirts have? If not A, even C will sell that. So if you have commercial alternative, suit for specific performance cannot come into picture. When commercial alternative is not available, is when I will demand for the product only. I don't want money. Getting it? Hello? Next one, suit for injunction. What do you mean injunction? Stay order. What is that? A and B, they are fighting over a land. They are in litigation now. There is a land dispute going on. Meanwhile, people, B started constructing one building over that land. Now, A goes to the court and says, sir, this dispute is going. How can he start building there? Can you please tell him to stop? Until this dispute is resolved, he cannot build anything. Now, the court passes one order. That order passed by the court is called as what? Stay order. In legal language, it's called as injunction. I can ask if someone is going ahead with the contract, I can go and get an injunction order, meaning stay order. I have that right. Here, hello? Next one, suit for quantum merit. What do you mean quantum merit? Now, for example, let us imagine if I come and teach you for 3 days, if my pay is say 1,000 rupees. Yes, sir. Now, if I have come 2 days, the last one day I was not able to come. Now, let us imagine the academy says we will not pay you even 1 rupee. Is it fair? Now, this is only called as what? Quantum merit. What do you mean by quantum merit? I have come for 2 days. Now, for that 2 days, whatever is my payment, that has to be given. Are you getting the point? This is called as what? Contract is divisible. Meaning 3 days, 1,000. I have come 2 days. I did not come 1 day. I am able to divide the contract. In such case, I deserve for the work I have performed. I have performed 2 days work and hence I will be paid for 2 days. Some contracts are indivisible. Example, sir, I have done 3 days class also. But after the class, you guys did not understand anything. You guys went and asked one more class. Sir, we want law to be done again, but by a different faculty. Now what happened? I have done my job, but I did not do it to the mark. Now, should Arivu give me 1,000 rupees only?
No.
Or can Arivu say we will give you 0?
Yes.
Now, this also is a case of quantum merit, where the contract is indivisible. Contract is completed. I cannot divide now, pay. Now what do we do? Now I need to appoint one more person. Now they might come and do a very small revision and he charged, let us imagine 500 rupees for it. Arivu can deduct that 500 from my pay and they will have to give me that 500 rupees at least. These are called as indivisible contracts. Example, another example, let us imagine I get this whole classroom painted. The person has come and he has painted the whole classroom, but the work is done shabby. Meaning it is clear, it is evident, he has messed it up. I need to get it rework done. Now he has done the work, entire day he has worked. I need to pay him some, say 2000 rupees for the work he has done. But there are patches. Now what do? I'll call one more person. I'll tell him to complete the work. For that, he charged me, let us imagine, some 500 rupees, 1000 rupees. Now, what I will do for the first person, I will have to make the payment. I will not say, because you have done a shabby work, I'll not pay you. I will make the payment, but I can deduct some reasonable amount for whatever I have to redo it. Then I can deduct it and I can pay the rest of it. Now, this concept is called as what? Quantum merit. As much as performed. How much ever I have performed, I deserve the payment for that. It cannot be a zero or it cannot be a full amount also. Understood? That is what is given here. If the contract is divisible, meaning 3 days, 2 day and 1 day, I can divide it. In that case, I can claim money for whatever I have performed. 2 days I can claim. Next one, when a contract is indivisible, what will happen? The party may deduct money for the bad work done, if any. Clear? Huh?
If the second faculty this contract is agreed to pay more than 1000, like first faculty is agreed to pay 1000. In that case, how it will be compensated?
It will actually go to ordinary damages. Now we will file a case saying that because of you, we incurred more cost. Now it will become a case of ordinary damages. So we can even expect some money from you if you have done such shabby work. Yes, sir. Okay, clear? Hello. Suit for injunctions. Okay, the last one, sir, suit for damages. Now, damages can be of various types. The first damage is called as general or ordinary. What do you mean by general or ordinary? What is general or ordinary? Whatever is direct cost, people, is called as ordinary damages. What do you mean by special damages? Special damages means, people, I have set certain special scenarios to you. I can recover the cost even for that as well. Example for general or ordinary damages, Hadley versus Baxendale. What is this general or ordinary damages? I mean, to tell it in a simple way, people, A agreed to sell 1000 shirts to B at a price of 1 lakh rupees for 1000 shirts. Now, because A did not deliver it, B rescinded the contract. B went and purchased the same shirts from C, same quality. But C sold it for 1.2 lakh. It's a clear cut. My cost has gone up by 20,000 because you did not perform. Agreed? If you had performed, my cost is 1. Because you did not perform, my cost is 1.2. Who will give me the 20,000? Under ordinary damages, I can claim 20,000 from A. Agreed? That's how ordinary damage. Hello? Pakana. Now, what do you mean by special damage? What is special damages?
I need that part. But during within specific time, I did not do, I can recover the whole amount. Yes.
Now, let us imagine this 1000 shirts. Why did B order from A? Because B got a very good order from probably some office. I had to deliver this 1000 as something like uniforms. Now, you did not deliver. Now, people, because of that, I lost around 3 lakh rupees because you did not deliver. Now, B filed a case on A. You need to pay not this 1 lakh. You need to pay me the 3 lakh rupees. Because of you, I suffered this loss. Now the question is A liable for this 3 lakh rupees which B lost because I did not supply? He was not able to deliver. For that, am I liable? Correct. The conditionals people, only one question is asked. A, B, did you tell this condition to A when you place the order? If answer is yes, then B can recover the entire 3 lakh rupees. If the answer is no, I did not tell it, I just placed the order, then you cannot recover this 3 lakh rupees. This is only called as what people? General damages, special damages. Special means what people? If you tell any special circumstances to the party, if you have conveyed it, then the party is responsible for the special damages as well. If the special damages are not communicated, the special scenarios are not communicated, you're always entitled only for ordinary damages and not for special damages. Clear? Yes, sir. Simple. Next one is vindictive or exemplary damage. What do you mean vindictive or exemplary? It is a matter of revenge. Generally, when will this scenario happen? See, when will this exist? It will happen when A promised to B that I will marry you. But A did not marry B. In such scenario, I can file a case, and that is only called as wherever, because it is emotional damage, it's a contract, you can claim. Yes, there's a case law also, Frost versus Knight. If you remember, that's a wedding scenario only. Frost versus Knight, you have no in your case. Yes or no? Next one is wrongful dishonor of customer's check. Always remember, people, there are two types. What is wrongful dishonor of a check? A gave a check to B, 1 lakh rupees. Go and deposit in the bank, you will get 1 lakh rupees. B came and deposited. A's account has money, but ICICI Bank says, no, sir, A's account does not have money. That's why they're telling you wrongful dishonor. There is money in the account, but they intimated that there is no money in the account. Now, because of that, in the industry, my reputation is gone. Tomorrow, if I give check, people will not believe. Now, I want to take revenge on ICICI. A will file a case on ICICI for vindictive or exemplary damage. Hello? Now, my question is, who is A? If A is a businessman, or if A is you and me, non-businessman. If it is a businessman, remember, people, by default, I need not prove anything. I need not prove that there was a damage. By default, I will get compensation. But if I'm a non-businessman, I'm talking about you and me. You and one check it, you know what happens in society. Who cares? Who knows? Correct? I don't know about you. Now, if my check is dishonored, who cares? You are all reputable people. Now I'm saying, now see, listen. Now, if at all, if it is non-businessman, now if our check is dishonored, we need to prove to the court what is the damage that we suffered because of this wrongful dishonor. If I can prove, even I will be entitled for compensation, but I need to prove. But a businessman need not prove. He will by default get compensation. Understood? Once they have asked this question. Clear? Okay, next one, nominal damage. What do you mean nominal? Amazon had to deliver you the product today, but they delivered you tomorrow morning. Macha, did you suffer any loss? Time is not essential, but did you suffer any loss? Nothing. But don't you think it's still a breach of contract? You can still file a case, no? Yes or no? Now, this is only called as what people? Nominal damage. Nominal means what people? Something which is small. Just to satisfy your ego, some damages will be given. It can be 100 rupees. If you actually look at Bare Act, it says, even it can be a 10 paise. Bare Act says. Yeah. So it can be even 1 rupee, it can be 10 rupee. I'm saying not 1 rupee, 10 rupee in reality, but it can be even say that 100 rupees. It is just to satisfy your ego. Yes, you won the case. For that, they will give you damages. That is only called as what? Nominal damages. Nominal damages, when will it happen, people? There is a breach of contract, but you have not suffered any loss. In that case, you will file nominal damages. Clear? Next one, deterioration caused by delay. What is it? Deterioration caused by delay? Deterioration caused by delay. For example, a farmer agreed to sell apples to a star hypermarket. Yeah, the apples had to reach on 1st Jan 26, but there is a delay in the transit. It did not reach on 1st Jan 26, it reached on 5th Jan 26. Because of that, the saleability of apples, the value has deteriorated. If I had sold on first, I might have sold it at 300 rupees per kg. Today, I will have to reduce it to 200 rupees per kg. If not, people will not buy because it is not fresh. Now, who will bear this risk? Technically, I said I'll give you an apple. I gave you an apple. I mean, that is delivered also. Who will bear the risk? That is only called as what? Deterioration during transit. I mean, deterioration caused by delay. Remember, if it's because we are speaking about deterioration, that means I'm speaking about some movable goods. Goods only, no, end of the day. It will be technically governed under Sale of Goods Act. You guys will see this again there also. Yes, sir. But yes, according to Indian Contract Act, what does it say? Damages can be recovered from the carrier. Who is the carrier? The delivery agents. It may be physical damage or it can be even loss of opportunity to sell. Physical damage is what? Apples literally broke. I cannot sell it. Loss of opportunity to sell means what? There is a reduce in value. 300 rupees apple has become 200 rupees apple. I can charge you for both. Clear? Last one is called as prefixed damages, also called as liquidated damages or penalty. Now, what do you mean by prefixed damages? Concentrate, concentrate. What is prefixed damages? A and B entered into a contract. A agreed to sell 1,000 shirts. In the contract, they both have agreed. If you do not deliver the shirt on time, if you do not make the payment on time, you will have to pay a compensation of 20,000 rupees for breach of contract. Where is it written? It is already written in the agreement you guys have entered. It is already written. If it is already agreed between the parties, we call these as what? Prefixed damages. Now, between us, if I do not deliver you the classes on time, what will you get? We have agreed, huh? We have agreed, huh? No, no, this is not prefixed damages. We will go to court. Court will order what is valid and what is sufficient. We will go as per that because we have not agreed anything. But in certain commercial contracts, they would have agreed. Now that is only called as what? Prefixed damages. If parties only have agreed, what will be the compensation? It is called prefixed. If parties have not agreed, then we will go with court's discretion. Whatever court thinks is right, they will order. Hello? Understood, huh? Now, sir, let us imagine two scenarios. Scenario number one, we have written, if I do not deliver shirts on time, I need to pay 20,000 as compensation. Scenario number two, if I do not deliver shirts on time, I need to pay 1 lakh as compensation. Same 1,000 material shirts only. 1,000, I mean, 1,000 quantity of shirts only. In one place, I have written 20,000. In one place, I have written 1 lakh. Value of the contract is same, 1 lakh only. Contract is for 1 lakh only. But in one place, we have agreed compensation as 20. In one place, we have agreed compensation as 1 lakh. Looking at 20,000, what will be your feeling? What will be your response? 20 only, no. It's okay. Even if I do not deliver, what is the maximum I need to pay? 20,000. It's okay. When you look at 1 lakh, how do you feel? Contract value is only 1 lakh. If you do not deliver, 1 lakh will be compensation you need to pay. Now, people, you will make the ends meet. You will work day and night. If laborers are not coming, you will become the labor. You will make sure that you will do the 1,000 shirts. Why? Because the value is like that. Correct? Huh? The intention of putting 1 lakh here is to create fear in you. The exam code you guys need to write is terrorum. Terrorum. Terrorism means what? The reason of including the word 1 lakh as compensation in your contract is to create that fear. Tomorrow, even one thought comes to you, I will cancel the contract. But 1 lakh should kill you. So it will make sure you will deliver the contract. Agreed? Huh? Yes or no? Then whenever that is the word, meaning if we are using it to create fear, we use the word called as penalty. Sir, 20,000, no fear and all, sir. We use the word called as, we have to distinguish, no. I cannot say 20,000 and 1 lakh. The words we use to distinguish. If it is 20,000, we call it as liquidated damages. If it is really a higher number, we call it as penalty. Clear? Huh? Now, if I ask you, how did you arrive at 20,000? There is a logical reason. Because in the market, if you are giving at 1 lakh, I will take another 5 quotations. The maximum I'm getting is 1.2 lakh. So there is a logical reason why I chose 20,000, because the next alternative person will sell it to me with a higher rate. That is 20,000. That's why I have charged 20. So there's a logical reason behind how did I arrive at 20,000. Because a competitor will charge 20,000. That's why I've arrived at 20,000. Now my question is, how did you arrive at 1 lakh? How? No reason, no calculation. It's a illogical calculation. It's a random number. There is no calculation involved when you are coming at penalty. Whereas if it is a liquidated damages, it is always calculated. It is not illogical, it is logical. That's the difference. Agreed? Huh? Now, sir, in India, there is no difference between the word penalty and liquidated damages. We don't differentiate all that. It is there in UK courts. Are you getting the point? Hello? Now, sir, let us imagine in the compensation, we have written it as 1 lakh. Now, A did not deliver the shirts to B. Now, B had to buy the shirts from Mr. C. How much did I incur? Let us imagine I had to pay 1.5 lakh rupees to buy the shirts. But in compensation, we have written that I need to pay 1 lakh. If I do not deliver, I have to pay 1 lakh. But how much extra did B actually pay? 50,000. Now, B has filed a case on A in the court that A did not deliver the shirts on time. So there is a breach of contract. According to the contract, he need to pay me 1 lakh rupees. So B is demanding 1 lakh rupees from A. Tell me, in Indian courts, what is the maximum money B will get? 1 lakh or 50,000? 1 lakh or 50,000? 1 lakh or 50? 50, sure. So remember, Indian courts will never order more compensation than what you have actually suffered. How much did you suffer? 50,000. Because we believe court is not a profit-making place. It's a justice-seeking place. Justice is 50,000, not 1 lakh. What did you suffer? 50. What I will give you is 50 only. Court is not there for making profit. Court is there only to give justice. Justice is 50,000. Agreed? No? Now let us imagine scenario number 2. I purchased the product from C, but this time it costed me 2.5 lakh. That is 1.5 lakh more than what B has, he would have got it from A. Now my cost has now gone up by 1.5 lakh. Now B has filed a compensation from A. I have asked for 1.5 lakh rupees. Tell me how much will I get? 1 lakh or 1.5 lakh? 1.5 lakh? 1 lakh. 1 lakh only, no? 1 lakh or 1.5? 1 or 1.5? The court will order how much, people? 1 point. How much will court order? 1 lakh. Why? Court will say, I would have given you 1.5 lakh. Why did you put an upper limit in the agreement? I would have given you, but you only said, sir, I would not want money more than 1 lakh. Where did you say? You have said in the agreement only. Hello, sir, to remember, easiest way, remember, always actual damages, meaning whatever you actually suffered or whatever is agreed in the contract, actual or agreed, whichever is less. In exam, if you get confused, then apply this logic, but don't write this in your exam. This whichever is less or all does not exist in your book. It is only for our ease of understanding we write. So it is always the court will order whatever you guys have agreed or actual compensation, whichever is less. Clear? Hello? Okay, that is your penalty and liquidated damages. Important, remember and go. That is your unit 5. Any doubts? Hello? Okay. Next one, sir. Unit 6, contingent contracts and quasi contracts. Okay. What is contingent contracts and quasi contract? What do you mean by contingent contract? Contingent means what? What is contingent? Contingent means what, people? An uncertain event. Something which may or may not happen is called as contingent contract. Contingent contract, there are examples of contingent contract. 2 contracts: indemnity contract, guarantee contracts. That's your next unit. Both are indemnity, I mean, both are contingent contracts only. But in short, what do you mean by contingent contract, people? A contract which is uncertain. Example is people insurance. You guys take a bike insurance every year. You have to take no insurance, bike insurance. Now, why do you take insurance, people? If I meet with an accident, then someone will give me money so that that money will not go from my pocket. Now, you tell me, pakka you will meet with an accident. I mean, that should know. But I'm saying, whoever has taken insurance, pakka they will meet with an accident. No, you cannot predict it. So, you will get the insurance money or not is uncertain. You may get it, you may not get it.
Conditions are needed.
Certain
Conditions to be followed. Insurance claim.
correct. Yes. No, I'm saying whether that event will happen or not, you never know. No.
Like if you go in triples, you get an accident.
No
compensation.
That is break of rule. Correct. That is also there. Yes. You need to follow terms and conditions. That is also there. But what I'm saying is, you never know whether on a normal day, whether you will meet with an accident or not. It's an uncertain event. You cannot predict it. Now, that's why such type of contracts are called as contingent contracts, which is uncertain. Agreed? Yes, sir. Regarding this, more will be seen in your next unit only. That is nothing but your indemnity contract, guarantee contract. One is the insurance, one is guarantee. Both we will see next unit only. Yes, sir. Hello. See, insurance, indemnity, guarantee. Both of it, that's your next unit only, no? Hello. We'll see that when we are doing indemnity and guarantee. Okay, rules regarding enforcement of contingent contracts. How do we enforce contingent contracts? How do we enforce? Meaning it is contingent. No, the Amazon and yours is certain. You know when to deliver, when to pay. Insurance, when does the insurance company has to make the payment? It's an uncertain event. So what is the moment when I can request for the money? When can I get the money from insurance company? So that is what they have given you. What is the rules regarding the enforcement of contingent contract? When can I get the money? They're telling you first one. It depends upon if the contract is for on an event happening. What do you mean by that? Now let us imagine on an event happening. Now there is a contingent contract itself on an event happening. Now what is this? Let us imagine A goes and purchase. Okay, let us imagine A wants to get some loan from ICICI Bank. Now ICICI Bank demands for some security, meaning some collateral. Now A will say, sir, I'll do one thing. I'll give you the collateral, But the collateral right now, I don't have it. Why? Because it is coming in a ship. I'm ordered for gold. I'm a gold merchant. The gold is coming in a ship. It will reach probably in 5 days. Once I get that, I will come and give you that gold. Meanwhile, can you please start the documentation process? ICICI Bank says, okay, your loan agreement, everything is signed, everything is kept ready. The only thing we are waiting for is this ship to reach and the gold should come. So what we are entering into? We are entering into a loan agreement. Now, when will I get a loan? I will get a loan provided something should happen. What? The gold has to be given to the bank. Now, people, that is only called as on an event happening. When can I enforce the contract? When will I get the loan? The moment I go and give the gold, that is when I can enforce the contract. Now, what if I don't give the gold? What will happen? The contract will come to an end. It's a void contract. Sir, what if while the ship is coming, something happens to the ship? There are high tides. The ship breaks, ship sinks. Now the gold also went down. Now tell me, what will happen to this loan contract? When entered, it was valid. Subsequently, something happened. It became invalid. Now what do I call this as? The contract becomes void contract because I know this cannot come to me anymore. It will not come. Agreed? Now, when the entire contract is dependent upon this event, you will get money if it happens. You will not get money if the event does not happen. So, for me to get the money, what should happen? The ship has to reach the shore safely. That is what is called as on an event happening. The contract is enforceable. That is, the loan agreement is enforceable if the ship reaches safely on an event happening safely. If the event does not happen, people, the contract becomes void. Clear? Sir, what if the ICICI Bank said, hey, what if you take 1 month, 2 months, 5 months to bring the gold? Let us have a fixed period. You have to come and give the gold. I know it is an uncertain event, but I'll give you 1 month time. I will wait up to 1 month. In 1 month, if you do not come, people, I will consider this contract as void. Now the ICICI Bank will wait for 1 month. If the gold does not come within 1 month, the contract again becomes void. The second rule of enforceability, event happening within fixed time. If it happens within 1 month, you will get the loan. The contract is valid. If it does not happen within 1 month, you will not get the loan. Hence, the contract is void. Hello? Now, sir, A worries. Sir, what if ship actually does not reach? So what will A do? A, to be safe, goes and purchases a insurance for this ship. Now you tell me, when will A get money from the insurance people? When ship does not reach, when the ship sinks, when the ship destroys. That is when he will get the money. That is the third rule of enforcement. On an event not happening, ship not reaching, I will get money. The first one, ship reaches, I will get money. Second one, ship does not reach, I will get money. Correct? Because that is how the contract is made. That is the third rule of enforceability. On an event not happening, it can be enforced when event becomes impossible. Like, what do you mean by that? If ship sinks, if ship breaks, if anything like that happens, I can go and demand my insurance money. Agreed? Hello? Sir, what if now our bike insurance, right? Now, if I take insurance today, will that insurance be valid for 10 years? Then it will always be valid for a specific time. All insurance contracts will come with a time. Remember that. Depends upon what insurance you are taking. If it's a bike insurance, the validity is 1 year. If you meet with an accident within this 1 year, you will get money. If you do not meet with an accident in this 1 year, after 1 year, if you meet with an accident, you will not get money. That is the next one. On event not happening within fixed time. Agreed? So within 1 month only, if this anything like this happens, I will be responsible. After that, I'm not responsible. So the insurance contracts, I am responsible if anything happens in this 1 year. After that, I'm not responsible. Agreed? So if ship does not return within 10 days or months is when I am liable. So if it is within fixed time, it should happen within that fixed time. If it is time is not prescribed, then it can happen anytime. Agreed? Yes, sir. Enforceability of contingent contract. Next one, on an impossible event. What if impossible event, people? Depends upon it is initial impossibility, subsequent impossibility. Initial impossibility is always void agreement. Subsequent impossibility is a void contract. Correct? Next one, upon conduct of a living person. I'll tell you when we are doing the Sale of Goods Act, this particular thing. Conduct of a living person. Yes, sir. Hello. Okay. Last one, sir, is called as quasi contract. What do you mean quasi contract? What do you mean the word quasi? The word quasi means people similar, resembles. Yeah. So the word quasi means people something similar to, resembles to. So quasi contract means something similar to or resembling a contract. Now, what do you mean by the word quasi contract? Nothing but people. In a normal contract, there will be offer, acceptance, consideration, all of that will be there. In a quasi contract, all that is not there. Offer is not there. Acceptance is not there. But still, it's a valid contract itself. Who is saying? Law is saying. There is no offer, there is no acceptance, but still it's a valid contract itself. Where, sir? Example, people. Best example is your wallet. Yesterday, you find a purse. Now, where is it written? Was there an offer or acceptance that you have to go and return it back to the owner? Is it anywhere you have agreed with the other party? Then why should you go and give back your purse? Why should you give back your wallet? Where is it written? That is only called as quasi contract, finder of lost goods. Law says it is your duty. Even though there is no offer, there is no acceptance, it is still a contract. You have to return it. Hello? Understanding? So finder of lost goods is a example. Next one, what else? What else is the example? First one, claim for necessaries. Agreed? So if someone pays money to minor for education, a person unsound mind or dependents upon them, I can claim the money back, provided it is limited to the estate. So if someone is giving money for minors education, it's not a contract, noda. Minors agreements are void agreements, but it is still enforceable. Quasi contract, clear? Okay. Next one, payment by interested person. What do you mean interested person? They'll ask you a question here. Quasi contract, you can expect a question. What do you mean payment by interested person? Now, for example, Arivu is staying in one building. It was clear that we will give, say for example, we will give 1 lakh rupee as rent to the landlord. The landlord has to take care of everything. That is rent, maintenance, electricity, water bill, everything is on him. Now every month we are giving 1 lakh rupees to the landlord. But let us imagine, people, the landlord has not paid the electricity bill to the the authorities. Now, because of that, the electricity department, the BESCOM department, they sent a notice to this building saying that if at all the electricity bill is not paid, we are going to take away the fuse and you guys cannot enjoy the electricity. Now, people, in spite of we giving here, we feared that, if at all they take away the fuse, our classes will be affected. And we paid the money to the electricity board. Technically, who should have paid? The owner has to pay. Then why did we pay? Because we also have some interest in this property. If at all he does not pay, I will also suffer. My revenue is also going. And that's why I am paying. Because even I have some interest in this property. Now, if I am making the payment, I made this 20K payment. The law is telling I have a right to recover it from the landowner. The question is there an agreement between us that if you pay, I will come and repay the money to you. Has he told us? No. But the law still gives us a right. If I pay it, I can later recover it from him under the grounds of quasi contract, which I did not have a right to pay. But even if I pay, I can recover it. Sir, what if he doesn't pay? Deduct it in the rent which you are giving. It is valid. And this is a quasi contract. Clear? Payment made by a interested person. Next one, person enjoying benefits of non-gratuitous act. What do you mean by this? Imagine you go to, what is that? You go to a hotel, service hall. You ordered for one dosa. Along with dosa, one vada also came. You started eating. When bill came, people, there is a bill for dosa and vada. Now you are saying, I ordered only dosa. Why are you billing me for vada also? Now you tell me, people, whether you have to pay the bill or not. You have ordered only dosa, but he has given you vada also. You ate. You have to pay. You can't go and argue there. Did I ask you to give? He will also ask you, did I ask you to eat? Because it is common sense in this world, people, nothing comes to you free of cost. Don't tell me Bobo is going, sir, buy one, get one free. So an offer is going on. Whatever. This is not the world. We all know there is nothing that comes to you free of cost. Yes, another question can come to you. For example, a person, while you're standing in a traffic signal, a person sprays the car spray, that is cleaner, the wind cleaner, the visor cleaner, and he starts cleaning, and you let him clean. After everything is done, he's coming and asking you some 20 rupees to be paid. 50, sorry, Damacha. 50 rupees he comes and asks you to pay. You tell me, should you pay or not? Should you pay? Sir, I thought complimentary. What? For standing in traffic signal. You know, in this world, nothing is free. You accepted the service. This can come under two. One is person enjoying benefits of non-gratuitous act. Second one, implied contract. Your acceptance is implied. You are allowed him to do. You should have stopped. Hello? By conduct only, no? They do it, no? They will start doing it. Yes or no? Okay. Last one is finder of lost goods. Should I give it a? If you find a purse, should you give back to the owner? He's saying, no, sir. You should give it, unfortunately. You are under a liability. It's your responsibility to give. Sir, what if I did not find the owner? You did not search only. Remember, people, it is your duty to search the owner. If you are not able to find it, people, then remember, whosoever found it will become the owner. You can use it until you find the owner. Clear? Hello? Holland versus Howler. A person. Now let us imagine, people. There is someone dropped probably their ring here. Yeah. So that person came and gave it to me. Sir, someone's ring, sir. I said, okay, I'll give it to the owner. So I said, people, there is a ring. If someone can prove it is yours with bill, with picture or something, then I'll give this ring to you. 5 days happened. We sent messages and all. We put it on YouTube and all. No one responded. Now, after 5 days, people, the person who found it, Nitish came and asked, sir, did you find the owner? I said, no, Nitish, I did not find the owner. Nitish is telling that, sir, give me back the ring. I said, Nitish, it is not yours. Why should I give it? He said, sir, you were not able to find the owner. Then give it back to the ring to me. Now you tell me, people, who should keep the ring? Nitish or I can keep it. I have spent money, I've spent effort, I've done YouTube video. I came and I draw the ring here. I said it is available. I took so much of effort. Now then, remember in law, whoever first found it will be the owner. Nitish will get a right to take the diamond ring, provided. Now, if I have spent some money, he must repay that expenses to me. Meaning, imagine if I have run some ads for that ring. For that, he has to pay for it. Correct, Noda? 10% I can keep. 10 na. You selfish fellow.
that book against the coins.
10% iರುತ್ತೆ. If the owner has to see, you will again see this in the next thing. What is that? Bailment, it will come. No, finder of lost goods. Now in bailment, you will see the continued version of this. Now imagine if I find the owner. Nitish found the owner. Now Nitish, to preserve this, he has spent some money. Now is the owner liable to pay that money to Nitish? Yes. Answer is yes. What if the owner does not pay that money? Nitish can keep the goods with him. But remember, Nitish does not have a right to sue the owner for the 600, 500, whatever he has spent. He cannot sue, but he has a right to keep the goods with him until the money is paid. Yes. Imagine if any reward was given. Someone has put a newspaper ad. If anyone who comes and gives me this ring, I'll give them a compensation of, reward of 5,000. Now it becomes a duty. If the owner does not give that 5,000 to Nitish, Nitish has a right to file a case on it, but not for the expenses. Only for reward you can file a case. Clear? Hello? Understood? Money paid by mistake or coercion. What is this money paid by mistake or coercion? You go and drink one tea instead of paying this. When now it is not happening. Initially, when our new notes came into picture, color, which color? Our minds are so used to, okay, this color means this. But in 2016-17, when that new notes came, pink, green, black, what and all came. Now, all of a sudden, green value people don't know. Now, if at all I've given some money by mistake, now I go to the shop, tea cost is say 10 rupees. I give 100 rupees by mistake. Now tell me, should the person give me back this 90 rupees? Now he will say, did I ask you to give? Why should I give? Correct, no. Offer irka, acceptance irka, but still contract irukku. That's why it's called as quasi-contracts. Understood? Law says it is your duty to return that. You all should come to the class then. Okay. Money paid by mistake or coercion. Done? Yes, sir. Okay. Done. Next one, Unit 7, Contract of Indemnity and Guarantee. Now, what is Contract of Indemnity and Guarantee? What is indemnity? What is Contract of Indemnity? Insurance is an example. Indemnity is nothing but
To make good the loss.
if someone promises you, if you suffer any loss, I will take care of that loss. Now, that is only called as people indemnity. A is a wholesaler. B is a, A is a manufacturer. B is a wholesaler. C is a retailer. Yes, now A tells B, I will supply you the goods. You further sell it to C. If you suffer any loss in this process, I will give you the money. Don't worry. So imagine B has agreed with lot of people to supply goods, but there is some delay in manufacturing. Because of that, B was not able to deliver goods to C. C filed case on B to recover damages because they are suffered loss. Agreed? Now, people, if A repays this money, this is only called as what? Indemnity contract. One of the example. What other example we can say? Insurance contract is also indemnity contract. ICICI, Lombard gives you an insurance saying that if at all your bike meets with an accident, we will give you the money. So indemnity contract means what? If you suffer the loss, I will make the loss good. I will make good the loss. I will pay the money for it. Such type of contracts are called as what? Indemnity contracts. Remember, life insurance can never be considered as an indemnity contract. Yes, life insurance can never be an indemnity contract. Why? If a person dies, what will you make good? Indemnity contract is simple. If you suffer any loss, I will make good that loss. How will you make good life? A person has died. Money is not making good their life. That's why life insurance can never be considered as an indemnity contract. It's an insurance only, but it is not indemnity. Clear? Hello? Okay. Contract of indemnity meaning a contract where one party promises to save other from any loss due to conduct of promisor himself or any other person. Promisor himself. A only did not supply goods to B. Because of that only B suffered loss. Next one is any other person, insurance, bike, someone came and hit, I am giving you money. So loss can happen from me only or from any other person. Parties of indemnity contract, indemnifier. Who is indemnifier? Insurance companies. Indemnity holder, you and me. Some special points. Mode of contract, it can be express or implied. Life insurance can never be considered as indemnity. It must fulfill all the essential elements of contract. Right of indemnity holder when sued. They have asked 2-3 times. Now, what is this? Right of indemnity holder when sued to recover from promisor. What do you mean by this? Rights of indemnity holder when sued to recover from promisor. A took an insurance from ICICI. A met with an accident. But ICICI did not make the payment. Now, A filed a case on ICICI because they did not make the payment as per the contract. Now, what and all A is entitled to? If you are directly paid, you have to pay only the accident cost. You did not pay it. That's why I came to court. Now, what and all A can recover? A can recover. First one, damages compelled to pay. What is damages compelled to pay? Damages compelled to pay is nothing but people. See, technically, I can get 3 things. One, whatever is the money as per the contract. Imagine if I have to get some 50,000 rupees for damages. I will get that 50,000. Correct? Okay. Now I came to court. Who will pay lawyer fee? Who will pay court fees? You should only pay. Add another 10,000 rupees. Sir, and main mental trauma. You know, no? Sir, how much? My God. All of this. Because of this, give me 1 lakh rupees. For Bisivadabad, mental trauma 65,000 they took. For insurance, it will be much more. Yeah. Okay. So I will get to what people. 1,60,000. Now this is what they said here. You can get the money, whatever the damages as per the suit. I'll get as per all sums paid under the terms of compromise and costs in defending the suit. One is I will get my contract amount. I will get extra damages amount. Damages is that 10,000. Sorry, 1 lakh. And whatever is the legal charges, 10,000 rupees. I'll get all these 3. Exam 2 times they've asked. Remember and go. Yes. Can happen. Why not? Recently there is one in YouTube also the case is there. Wife, you know this divorce case, no? Wife has asked as a maintenance alimony. Wife has asked 6.5 lakh rupees for maintenance per month. 6.5 lakh rupees. It's there. It's the entire case. 6.5 lakh maintenance case you put. It is there on YouTube. You'll get that. Correct, correct. Yes. It's a lady judge only, that too. Lady judge. She says, all these frivolous claims and all, I cannot entertain. A person, why does they need 6.5 lakh for a living? The concept of maintenance and alimony was to make sure you get support. If you want 6.5 lakh, the lawyer would have come on behalf of the client. They will tell, the judge tells to the lawyer, tell your client to go and work and earn the 6.5 lakh rather than exploiting from someone. See, 6.5 lakh they have asked. It happens. Yes, all that happens. Such cases happen. Mental trauma and all will always be there. Yeah. Contract of guarantee. What do you mean guarantee, pa? Guarantee. A, B, C. Correct, huh? A takes loan from B. What is A's name?
Principal return.
You will call A as principal debtor. Whoever gives loan, what do you call them as? Whoever gives a. If A has taken 2 lakh rupees loan. If A does not repay, C will repay the loan. What is C called as? Surety. How many contracts are there in contract of guarantee? This is the first contract, the contract between principal debtor and creditor. This is called primary contract. There is a second contract. The secondary contract is between whom? The surety and the creditor. There is a third contract. That is between whom? The principal debtor and the surety. This is only called as what? Implied contract. That means what? Hey, if you do not pay 2 lakh, I will have to pay. So if A did not pay, C paid on behalf of A. Technically, why should I suffer loss? The law gives me a right. Okay, today I will pay, but tomorrow I will recover it from you. Law gives me that right. It's an implied contract between these two people. That if I give money on your behalf, someday you need to repay it to me. That's the third contract. Hello. Understood? So, if C has paid money on behalf of A, now C has a right to recover the money just like a creditor. Whatever rights B had, same rights C will have. Hello. What is this process called as? Subrogation. Very good. What if C is liable only for 1 lakh? That only I can recover from here.
How we can recover from see the
See, if B needs to get 1 lakh rupees.
like A got loan from B like 2 lakhs.
Huh.
C is only to give for 1 lakh.
Huh.
A didn't able to pay 2 lakhs.
Huh.
Like B, how C
Okay. So you're saying that 2 lakh is the loan amount, but surety was only for 1 lakh. Now, next question is, do you have any security? Generally, in your case, whenever half is only security, the half will be surety. So there will be some gold or something involved. Let us imagine nothing is there. Then it's always a loss of 1 lakh. You will not take it from the surety. Yes, sir. Okay, surety, principal, creditor, done. There are 3 contracts, principal, second, implied, done. Okay, done. Next one, essential features of a guarantee contract. What are the features done? First one, there has to be, for a guarantee contract to exist, what is important? There has to be a principal debt. Agreed, huh? Tell me people, in these 3 parties, who and all can be minors? Can A be a minor? A be a minor? The borrower, principal debtor, can he be a minor? Definitely possible. How can minor be? Can A be a minor? Yes, sir, A can be a minor. Minor agreements, rule of minor agreements. He can be a beneficiary. Incoming okay, outcoming illa. Yes, sir. So incoming is okay. You're a beneficiary, allowed. Yes or no? And there only you saw, whenever there is a contract where the minor has borrowed money, if surety is a major, surety will be liable. Now tell me, can a surety be a minor? What? Consideration, guarantee without consideration is void. Of course, consideration should be there. That is a loan. But no need of any direct consideration between surety and creditor. Of course, between us, it's not there. On behalf of me, borrower is taking. Principal debtor incompetent, surety incompetent cannot happen. Existence of liability, it must be enforceable and not a time barred debt. Meaning, surety when he is giving a guarantee, that time the loan should have not become time barred. Only then it will be valid. That is, the 3 years period should have not been over yet. Yes or no? No misrepresentation or concealment. What do you mean by this? No misrepresentation or concealment.
Terms and conditions between the participating.
So I had one student. The student sent me an email. Sir, if you don't mind, I need a reference letter from you. I said, why? Sir, in my office, it's a procedure that we have to take a reference letter from some people. So one student asked, sir, can you give me a reference letter? Now imagine people in a good faith. What do I know? Okay, student only. So I will say, okay, I will give you the reference letter. Now, what do you mean by this representation or concealment? Now, I don't know why this reference letter is asked. Now, imagine the reference letter is being asked because this person, in the place wherever this person was working, this person has done some fraud. What fraud? Embezzlement of cash. What embezzlement? Inflation of bills. Meaning what? If I go and come in a cab, 200 rupees, no. Isa, 300. Embezzlement of cash. Now, certifying his character, after 1-2 months, they're asking if you want to continue, you have to get some certificate from any of your, say for example, any person, working professional, you have to get a reference. Now, my question, did their firm, let us imagine it was a CA firm, did they give me this background? Answer is no. They just asked me for a reference letter. We gave a reference letter. Now, people, it is your duty to tell as a creditor or any person, it is your duty to communicate why this particular reference is being asked for. If you are concealing the facts, you did not tell me that this person has already done all of that, then I wouldn't have given. If you conceal these facts and take a guarantee from me, my right is not affected. I will not be liable for any of his mistakes. My surety right will come to an end. I will not be liable. That is what is this. No misrepresentation or concealment. Any guarantee obtained by creditor by silence or misrepresentation shall be invalid. Clear? Yes, sir. Next one. Need not be in writing. Oral is also valid. Of course, Indian Contract Act. Guarantee is not valid until court is imposed by surety. What do you mean by this? A and B. B is asking for a surety. What is the value of the loan? 10 lakh. A came and said, hey, Mr. Say, for example, D, can you give me a guarantee for this loan? D said, I will give, but one person alone, I can't handle 10 lakh. I want at least another 2 more people. What I can maximum give is 3 lakh. I want at least another 2 more people. If not, mine also is invalid. If I have clearly put this condition, I'm saying I'm liable for 3 lakh. That too provided. If there are other co-sureties, if I have clearly said this communication, then people, I am not liable until co-sureties join. Let it be even for the 3 lakh. I will not be liable until the co-sureties join. That is what is this condition. See, guarantee is not valid until some other person joins as co-surety if such condition is imposed by surety. Clear? Hello? Understood? Okay, types of guarantee. Specific guarantee, continuing guarantee. What is specific guarantee? A took one loan, 1 lakh rupees. For this loan alone, C gave a guarantee. It's called as specific guarantee. A is taking loan from B, business loan, OD facility. I might be taking loan in 1 year. How many ever times is possible? Now C will come and tell, okay, I'm giving a guarantee for a period of 1 year. In this 1 year, whatever transactions A do, I will be liable. So a guarantee which will extend to series of transactions, not for one. It can be 3, 5, 10. Such type of guarantee is called as what? Continuing guarantee. Can I revoke the continuing guarantee? Very good. Past transactions can never be revoked. Future transactions can be revoked. And remember, upon death, automatically all the future transactions will automatically be revoked. Sir, what do I mean by that? I gave a guarantee on 1st Jan 2026. I said it will be valid till 31st December 26. I want to revoke it on 1st June 26. Anything happened in the past, I cannot revoke it. Anything that is going to happen in the future, I can revoke it. A continuing guarantee, I cannot revoke the past transactions. I can revoke the future transaction. Exam they have asked. Clear? Huh? Hello? Okay. Nature and extent of surety is liability. Liability of surety is coextensive. What do you mean by that? Exam, they can ask you. Coextensive means what? Sir, loan is 1 lakh. Interest on the loan is at 10% per annum. That is, I need to pay 10,000. The surety's liability will be 1.1 lakh. Whatever is principal debtor's liability, surety liability will be same. Sir, what if in this 1 lakh, the principal debtor has paid 40,000, 60,000 is remaining. Coextensive, whatever he needs to pay, my liability will be same. Hello? Done. Liability of surety is secondary in nature. Agreed? That is only if principal debtor fails, the surety will be liable. Hello? People, let us imagine a loan had to be given. The loan had to be repaid on 1st January 2026. On 1st January 2026, the principal debtor did not repay the loan. The creditor directly filed a case on the surety to recovering the money. The surety is telling, hey, the time period is over, but you cannot directly file a case on me. You have to first file it on principal debtor. But the creditor directly filed a case on the surety to recover the money. They have come to you asking your opinion. Is this valid? Can I direct? So can I directly file a case on surety? Is it valid? Yes or no? Yes, people, I can file. What is the date of repayment? 1st January 2026 the date of repayment. Did you pay? No. If at all on the due date, if the money is not paid, I need not first file with principal debtor and then come to surety. I have a direct right to come and file a case on surety. Exam question, no. 100% wrong answer. Liability arises immediately on default by principal debtor. Hello? Okay, defect in document. Debtor and surety both are discharged. Remember, unenforceable contracts. Based on validity, types of contracts. Any contracts which have technical errors, spelling mistakes, I cannot bind the principal debtor. Even surety is also not liable. Creditor can sue surety directly. On the last date, not in between. On the last day, if it is not paid, I can directly go. Clear? Okay, next one. Discharge of surety. When will surety be discharged? First one, by revocation. When will the revocation happen? First one is notice. I will clearly say, sir, I have given 1 year. No, I want to take it back. Always you can take back. Past, you are liable. Death of surety, what will happen? Question no. They will ask you here. Future transactions, if it is a continuing guarantee, if there is a death of surety, future transactions will be revoked. What about the past transactions? His property will be liable. Whatever is the value of the property, that will be liable for the past transactions. Remember that. Next one, by novation. What is novation? We already seen if there is a change of contract, of course, the parties are discharged. Old contract replaced by new contract. By conduct of creditor, variance in contract without surety's consent. What do you mean by that? A has taken loan from ICICI Bank. The loan agreement was 2 lakh rupees. For this, I've given a surety. C has given a surety. But people, they have now not made the loan for 2 lakh. They have increased it to 4 lakh. There is variation in the terms of the contract and the C is not aware of it. C is discharged. So the rate of interest was 10 percentage. Now it is being made 14 percentage. Is C aware of it? No. If you're changing any terms without surety's knowledge, surety is discharged. Hello. By release or discharge of principal debtor, enters into fresh contract with principal debtor, does any act or omission. What do you mean by this? ICICI Bank is say, hey, yeah, you goda, I'll not do anything to you. I will directly go and catch C. If you're releasing him, he is also released. Agreed, huh? That is what they have given you. By release or discharge, enters into a fresh contract with the principal debtor. There is the first contract. For technically it comes under novation only. There is one more contract entered. Then of course I'm not liable for that. That is what they are trying to tell you. For example, we are all going behind Vijay Mallya, no? Vijay Mallya. Hey, Vijay Mallya is liable, ada. Vijay, Anna podcast no. Huh? Vijay Mallya is not liable, ada. He told like that, sir. Vijay Mallya liable or not? Vijay Mallya is liable. Vijay Mallya is liable. Then what did you see in that podcast? First of all, people, Vijay Mallya never borrowed the loan. Who borrowed? Kingfisher Airlines borrowed the loan. Correct. So now tell me, is Vijay Mallya? Now that case, why am I telling here? There should be something else, no? What is the topic? Macha, remember, why we are behind Vijay Mallya is because Anna was the surety for the loan taken by Kingfisher. Understood, That is why we are behind Anna. Recently, now, as you guys would have seen in that podcast, there were 3 sureties, including one of it, Reliance. ಆಮೇಲೆ ಟಾಟಾ ಇನ್ನೊಬ್ಬರು ಹಾಕ್ಬೇಡ Vijay Mallya, and it was all companies. United Breweries was one of it. That's why they are all now behind them. So technically, as per the recent verdict, 14,000 crore worth money has been recovered from Vijay Mallya. That's why he's saying if money is repaid, then why are you still against me? You know what? First thing that happened to him, he went to UK, no? Indian government seized Vijay Mallya's passport. So Vijay Mallya cannot travel anywhere. Without passport, how will you travel? That's why who cares? Even if money is there, he's not able to leave the country where he is in. That's the first thing that they did. And what is the total money that Vijay Mallya had to pay? Something around 8,000 odd crore, around 9,000 crores. 6,000 is loan amount. Along with the interest is around. For example, yesterday only there was one income tax. One person had come for some opinion. In 2014-15, some transaction has happened. The value, they are saying that they had to pay a tax of around 97 lakhs. He has got a claim notice now, 2014 transaction. So he should have paid IT of around 97 lakh in 2014. He has not paid. In 2025, he has got a notice. That means 10 years has elapsed. Correct, no? If you had paid that day, it was 97. You have not paid till then. That's why he has to pay interest now. He interest is come to 37 lakhs. Plus 97 lakhs. So I'm telling, but there is time. IT people cannot go beyond 8 years. That's the maximum time. But in this case, they have already initiated a proceeding somewhere in 2020. This was a reminder notice. And this person is an NRI. So in 2024, when he had come to India, that is when he got to know, okay, all this has happened. See, now second question number 2. IT notice has sent. He did not receive it because he is not in India. He's saying, I was not aware of it. Is it a valid excuse? Mistake of Indian law, valid contract. You need to pay. No excuse. You have to pay interest. You don't have a choice. You tell 500 stories. I'll tell you my case only. Listen, I'll tell you. I'd been to one place. It's called Vietnam. So I'd gone there. I had rented a bike. We are all used to driving left and right, right? So in Vietnam, it's opposite. Our mind is so used to it. I took a left turn where I had to take right turn. Anna, Allah stopped. What will I say, sir? I don't know. Did he leave me? Answer is no. He levied me $50 penalty. ಮತ್ತೆ ಕಟ್ಬಿಟ್ಟು ಬಂದಿಲ್ವಾ then you have to pay. Mistake of foreign law, for them it is their law. Correct pa, when you are in the law of their land. In MDH case, you are in India, they are in foreign. There is a contract for the goods. Here I am not goods, I am there. So when I am there, I have to follow their land. I know Bharat Mata ki jai, but there I can't. I had to pay. First of all, they don't understand our language. English is like around 5% of the people can speak. Full trip will be like this only. Google Translate, Rana. See. Rana, I was like, hey, he is not getting, he is not understanding. This Google, I don't know what it is translating. I know I believe Google, but only to one extent I can believe. Then what can we do? You have to pay. Same thing applies here also. He is an NRI, but you belong here. Mistake of law can never be excused. You have to pay. Yes. No, Vijay Mallya, why is he liable? Is because in the capacity of a surety. The entire chapter is him only. Anna. See, at times surety. Did he think Kingfisher Airlines will not be able to pay? If he had thought, why will he give his personal asset as guarantee? 14,000 crores. One not two. For $50 only, even now I wake up in my dreams. Oh, imagine 14,000 crores. What will be the effect? ನಿದ್ದೆನೇ ಬರಲ್ಲ. So that is how it is. That's what I'm saying. So it depends. Agreed? ಏನೋ ನಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾಗ್ಬಿಡೋದು. Okay. Okay. So enters into any fresh contract, novation, I told you. Does any act or omission legal consequences discharge of principal debtor? You do anything. If principal debtor is discharged, even the surety is also discharged. Second one, sir, by conduct of creditor. What are we seeing? We're seeing discharge of surety. When and all the surety will be discharged. If the creditor compounds, compound means what? Compound. Compound is nothing but compromise. Banks had to get 9,000 crores from Vijay Mallya. If imagine banks had, Kingfisher Airlines, if banks had entered into any compromise with Kingfisher Airlines, Vijay Mallya would have been discharged. Compromise means that if you guys enter into a contract, I am discharged. You guys agree something privately, I am discharged. Agreed? Okay. Gives time. Sir, 2 years is the repayment. I'll give you 5 years take. Surety is also discharged. Third one, agrees not to sue principal debtor. Bank is telling I will not file a case on Kingfisher Airlines. I will file on Vijay Mallya only.
What if Vijay Mallya dies?
What if?
Vijay Mallya dies.
Assets.
What if he does not have restricted property?
Why? Oh. ಇರುಕಾ ಇರುಕು ಏನ್ ಸರ್ ಅದು ಹೂವ ಏನೋ ಅಂದಿ ಕಿರ್ಚಿದ್ರಿ ಆರ್ ಸಿ ಬಿಡಾ ಆರ್ ಸಿ ಬಿ ಬುಳಿಕ್ ಆರ್ ಸಿ ಬಿಡಾ ಒನ್ ಆಫ್ ದ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ನೋ United Breweries and all these ways your assets only, no? Anna had one building da, that building went for an auction of 1,400 crores. Ah, this one da, UBC. See da, lived life king size. Anna actually lived. Hey, 20 floor building da, upon that imagine one mansion da. Ah. Literal bungalow. I think you guys would have seen.
Yes, sir. That symbol is still there.
It's still there. I mean, it's there. You just search UB City. It's there. He has a mansion on UB City. Okay. Next one, sir. Creditors act or omission impairs surety's eventual remedy. Macha, what is this here? Exam, they've asked. Creditors act or omission impairs surety's eventual remedy. A has taken loan 2 lakh from ICICI Bank by giving gold as security, and he has also taken surety from C. Now, the bank's negligence, they lost this gold worth almost 1 lakh, and A did not repay the loan. 2 lakhs is not repaid. Now they have filed a case on C to repay 2 lakh rupees. You tell me how much should C repay? Why? Now read. Creditors act or omission. Who is creditor? ICICI. Your act impairs surety's eventual remedy. Impairs means what? If you had kept this gold safe, my liability would have been reduced by 1 lakh. Because of you, my liability is now coming to 2 lakh. It is because of you. Then you only bear the risk. My liability will reduce by the amount of that security. So in the 2 lakh, the 1 lakh, whatever you lost, my liability will be 1 lakh only. Clear? Huh? Hello? Next one. By invalidation of contract of guarantee. When else it will be discharged? When the contract of guarantee is invalidated. When will it happen? First, guarantee was obtained by misrepresentation or concealment. Reference letter. Sureties come to an end. Contract that creditor shall not act until co-surety joins. Vijay Mallya said, I want at least another 4 more people. If there is no other people, then I am also not liable. Co-surety should join if a condition is there. Here, hello. Last one, sir. Rights of a surety. First one, against principal debtor, right of subrogation, which we have already done. If I pay the money on your behalf, I have the money to recover from you. Correct? Huh? Next one, implied promise to indemnify surety. Nothing but if I pay the money, there is an implied contract. You have to pay for it. That's the right against the principal debtor that the surety has. Agreed? Huh? Next one, against the creditor. What are the rights the surety has? Right to benefit of. What is this? If principal debtor has given any security, gold, in the previous case, even I have a right over it. Next one, right to set off. Sir, principal debtor has paid 50,000 out of the 2 lakh debt. Now, how much should I pay? Why? How did you say 1,50,000? He has already paid. No, that only is called set off. If he has paid anything, my liability will be set off against that. Right to share reduction. What do you mean by that? A has taken 2 lakh loan. A become an insolvent. A has assets worth 40,000 rupees. It is not given as security, but he has assets worth 40,000 rupees, and the bank recovered that 40,000 worth assets. Then the surety's liability reduces by that 40,000. I am liable only for 1.6 lakhs. That is the meaning of right to share reduction when principal debtor becomes insolvent. I hope it is clear. Hello. Next one, right against co-surety. What is that? They are liable to contribute equally unless otherwise agreed. Co-sureties having different sums liable. Important. I hope you guys know. This is easy, da. Okay, A has taken 6 lakh loan from B. Who is the surety? Surety is the C, D, E. C has given a surety for 3 lakh. Now, let us imagine A has paid 1 lakh. 5 lakh he has not paid. Now, how will you share that 5 lakh between C, D, and E? 1, 2, 2. Who has to pay 1? E has to pay 1, 2, 2. Agreed, huh? So let us imagine scenario number 2. A paid 4 lakhs. How will you share the liability? 2 lakh is to be paid. How will you share it? Simple, da. 2 lakh divided by 3. Equally, no? No. Okay, tell how much. Tell me how much.
Give the sureties, like say give 3 lakhs now, sir. See, first you have to give 3 lakhs.
Okay, so first 2 lakhs, whatever, you take it from C. Whoever gave the first surety, you take money from him. Next to from
C gave 3 lakhs now, sir. First C gave surety, so we have to first start with C, then from D.
and then from E.
And 75 and 50.
75, 75, 50. Okay, any other answer?
310.
310. Okay, anyone? Any other answer? Equally.
No, sir, not equal.
Any other answer? Four, 1, 2. Day liability only is 2 lakh. Da.
1,60,000, 30,000.
Yeah.
1,60,000, 30,000.
1 lakh 60, 30, 30. Day one question. 5 answers I got already. 1 lakh 60, 30, 10,000. Take something from him also.
10,000 should be D and E. D and E. 65 and 35.
Remember, people. 1 lakh 55. 1 lakh 50, 50.
1 lakh 65,000, 25,000.
1 lakh 20, 1 lakh 50, 25,000.
1 lakh 50,000, 25,000.
Where is this poor surety coming from? Da? You are paying a 25,000. Da. Yeah. 8 answers. So. People, answer is 2 lakh divided by 3. That's all. Remember, people, never take the answer in ratio. Hey, how will you take it? I have said 3 lakh. You have said 2 lakh. He has said 1 lakh. Now, just because the liability is coming to 2 lakh, you are saying take maximum from C. Why? Who says that? Why recover maximum from me? So remember, as much as possible, it is your duty to recover it equally. If it is not possible to recover it equally, then you recover it in a proportion. Now, what do I mean by that? Now, for example, let us imagine I have to recover 2 lakh. Share it amongst everyone. Why one person has to pay less, one person has to pay more? So for 2 lakh, it will be divided by 3. That's the answer, whatever you're getting. Okay, let us imagine if 3 lakh I need to pay. How will you divide it? Now everyone can afford it. So share it equally. Wherever possible, how much ever is possible, you have to share it equally. So 3 lakh again will be divided by 3. Because what? His liability is 1 lakh. He can take up to 1 lakh. Up to 1 lakh, share it equally. Now tell me, 4 lakh, how will I divide?
3 lakh 3 into 1 lakh.
See, up to 1 lakh, I can divide equally. Yeah. Now, after this, E cannot come into picture. Now, 50,000 is left. Now, see, this fellow is liable up to 2. This fellow is liable up to 3. 50, 50. Put it here. Equally. How much ever possible, you have to divide it equally. Just because one person agreed to pay more money, you cannot recover everything from him.
These are not like he gave first surety, so
Oh, you mix that appropriation of payment. FIFO. Okay, now tell me 5 lakh. How will you divide?
3 lakh
3 lakh?
first 3 lakh.
Macha, this is how you need to write in your exam also if it coming up. For our understanding, first to take who has the least payment. Up to that extent, you have to divide. So 1 lakh is the least payment, correct? Now still 2 lakh is there.
1 lakh.
Correct? Now I can divide it because this fellow's next is 2 lakh. That's the next least payment. Put another 1 lakh here. Now next scenario, 6 lakh will come here. Understood? That's what. Correct? That's how your liability happens. Directly I answered first only, much equally. After that you guys gave answers. No, that's the brilliance. After that you gave 8 answers. Okay, done. Yes, sir. Remember, exam point of view, they can ask a question here. Important. And it has been asked 4 times, sir. And wonderful thing is, every time they'll answer wrong. Love you, Dakanna. I know you believe in right to equality. Okay. You want a 10 minutes break? Yes, sir. Break the चाहिए. ये सब किसको चाहिए? Go and come. Okay, unit 8 people. Let us start with bailment and pledge. Okay, what do you mean by bailment, people? Bailment is nothing but a temporary transfer of possession. Possession of goods from one person to another person. Once the purpose is achieved, the possession will be transferred back. It's called as bailment. Ownership will be with you, only the possession will be transferred. Remember, if ownership is also given, it becomes a sale. So only the possession of the goods is given, it becomes a bailment. Bailment can be of 2 types. One is bailment without money, bailment with money. That is only called as gratuitous bailment, non-gratuitous bailment. Gratuitous means free. Non-gratuitous means not for free, meaning money is involved. Any example for gratuitous bailment? Giving a book to your friend is called as a gratuitous bailment. You're not expecting money out of it. Non-gratuitous bailment is nothing but you renting a bike, Zoom car. The ownership is with Zoom. You are enjoying the possession of the goods. It's a non-gratuitous. You are paying the rent for it. That is called as what people? Non-gratuitous bailment. Yes, sir. If you guys remember, under exceptions to quid pro quo, you have seen bailment will come there. Why it is coming? Because of gratuitous bailment. Your notes, your friend borrowing your notes, you are not giving money for it. But still it's a valid contract. That's why it is coming under exceptions to quid pro quo under unit 2. Clear? Okay. Parties of bailment, 2 parties. One is called bailer, bailee. Bailer is a person who gives the goods, the owner of the goods basically, or the person who transfers the possession. Bailee is the person who is receiving the possession. Essential elements of a bailment: contract, it can be express or implied. Delivery of goods, remember it can be only movable. Actual delivery, constructed delivery, anything can happen. Purpose, people, it can be for a particular purpose. After that, you will transfer it back. Example, my mobile had to be repaired. The purpose is repair here. After the repair is done, I will get back my mobile.
Possession having just custody is different from possession. You can expect a question. What is the difference between custody and possession? Is it different? So, for example, Nitish has gold. Nitish takes all this gold. He opens one locker in a bank. He deposits all that gold with that bank. He locks it. He brings back the key. Now, Nitish's gold is in SBI. Now, this contract is called as what? Is it a bailment or not? Is it not a bailment? His gold is with SBI now. Is it a bailment or not? It's not a bailment? Yes or no? It cannot be called as a bailment because people, what SBI has is just a custody and not possession. What is the difference between the word custody and possession? Custody is people, you're having someone goods with you, but you have no control over it. Custody, you have someone's goods with you, but you have no control over it whatsoever. It's called custody. Possession means people, you have someone goods with you, but you have some control over it. You take Zoom cars, it is under your control. You go right, it will go right. You go left, it will go left. Now, SBI, can they shift the locker from one place to another place? Can they check how much gold is there? Do they even know what is there? Though it is the locker in their premises, they don't even know what you have kept there. Our Indian movies, correct? No, Tata would have kept some secret map there. That's where the adventure starts. Correct, Noda? Now, the bankers do not know what is there in that. Another best example, what? Harry Potter movie, you guys have seen. Full gold. That is called as what? That is called as this only. It's a custody. They don't know what is inside. That's the difference. Clear? Possession, you have control. Custody, you don't have control. Clear? Okay. Now, once the purpose is done, you will return the goods. Bailment can be two types, gratuitous, non-gratuitous. Rights of a bailer. What are the rights of a bailer? To terminate the bailment. Bailer means what? A person who is giving the goods. What is his rights? To terminate the bailment. If bailee acted inconsistent with the terms of the contract. Meaning what? I've taken Zoom cars for 1 week rent. I've taken Zoom car for 1 week rent. Can I terminate the contract? Yes. They are telling you I can terminate, provided if I'm using the goods inconsistent with the terms of the contract. Inconsistent means what? I took it for within city transport, but I'm taking the car to Chennai. We are going it beyond the state. Technically, I'm not supposed to. That is the agreement we signed. Now, if I'm acting inconsistent with the goods, then people, they have a right to come and terminate it. They will not wait for third day. Imagine there is a speed limit. You're trying to exceed that. They have a right to come and terminate the contract. If you're doing inconsistent, they will terminate the contract. You're taking Paramatma and driving. Next one, premature termination. Premature termination, remember, there are two types of bailment. One is free, one is for rent. Meaning one is for money, one is free. Premature termination cannot happen in a bailment which is for money. If you want to do premature termination, it is possible only when there is inconsistent use of the goods. That is, I have taken Zoom cars for 1 week rent. Can they come and terminate the contract on third day? On a normal day, they cannot terminate it on a third day. But if they want to terminate, then it has to be only grounded inconsistent use of the goods. So the other type of bailment, your friend has given you the notes to copy and they have said it's okay that you take 7 days time. But on third day, they call you and say, I want my notes back. Can they demand it? Demand it, they can slap and take it from you. Free, on free, you don't get any right. They can demand it, they can take it whenever they want. Hello. Pakana. But remember, if at all you took the goods, let us imagine there is now Nitish is there, Jiva is there. Jiva is there. Jiva is no longer there. I mean, the class done. That's, yeah, you and your okay. Now, people, one second. Premature termination. Okay. Something. Okay. Understood. Idu. Yeah, okay. Jeeva and Nitish. Now, people, Nitish has one TT, tempo traveler. Yes, unused, lying in his garage. Now, Jeeva says, Macha, give me the TT. Jeeva Tukti. I will like to it. Give me that TT. Now, people, Jeeva came and asked, if you're not using it, can you give it to me? He said, how long you want? You give it to me for 2 years. Is it okay? He said, okay, take the matcha. Anyways, I'm not using it. Now, did he charge anything? Answer is no. He did not charge. Now, this TT was lifeless. No Jeeva. Now, people, what did Jeeva had to do? Jeeva had to take that TT, clearly wash it, paint it, tires had to be changed, revamp it. All that he put a lot of money into it. He at least spent some 40,000-50,000. After doing all of that, it's been just 20 days. Now, Nitish Anna came and said, hey, Jeeva, give me back my TT. Now, people, he's asking back his TT. Now, the question is, was it a gratuitous bailment, not gratuitous bailment? It was for free. I did not even charge 1 rupee. It's a gratuitous bailment. According to the rule, gratuitous bailment, I can come and cancel it whenever I want. Agreed? Now, he's coming and asking back. He said 2 years. He's asking back in 1 month. Now, whether Nitish will get back the TT or not, he will get it, provided the law says one thing. If at all Jeeva suffers any damages because of this premature termination, remember, Nitish, it is your liability to pay for that compensation. He cleaned it. He had to do all of that. Now, for that, you need to pay. He had to repaint it. You need to pay. Because on your word, he has done all of that. Now, this is only called as what people need to compensate bailey in case of loss. Simple, huh? Next one, suit against wrongdoer. TT was going. TT hit someone. Now, who can file a case? Remember, Jeeva also can file. Nitish also can file. Bailey can file. If there is an accident that has happened, who will file a case? Jeeva also. Bailey also can file. Even Nitish also can file. Anyone has a right. If a third person does any injury to goods in possession of bailey, bailer may file a suit against such person. Bailer means what? Nitish. Nitish also has a right. Clear? Huh? Right to sue the bailey. Who is bailey? The person receiving. What rights I have against the bailey? I can file a case itself. When compensation for loss by negligence of bailey. I have given TT. Anna bond has literally, there is too much of damages to the TT that is made. I can file a case for compensation allowed. Next one, compensation for unauthorized mixing of goods. What is unauthorized mixing of goods? Imagine my goods are also there. I mix your goods also with my goods. In such case, people, I will be liable to repay the money for the mixing of goods. In your exams, something and all, they'll ask the nonsense questions and all, they'll come. For example, A, B. B had one 10 kg of rice. A was not at home. That's why A had ordered rice bag at that time only. That rice, because A is not there, the delivery Anna will deliver it to B. Now the rice bag will be with B. Now B's son, useless fellow, will come. He will open the bag. He will mix this rice and that rice. So now it is mixed. Who will bear the risk? Exam question. Something and all they'll ask. But yes, that's a question only. Actual question only. Who will bear the risk? So answer is simple. If you can separate it, I know you have talent. Issa karka issa, gali mein issa you can do it. Correct? No. Turn on fan. Ille. Issa marka issa. Separate. It'll happen. No. No. If you are so talented to separate it and give it back, we know we are not talented. Pay the compensation. That is what they're telling you. Clear, huh? But we have to appreciate for the person who made this question. That too, I like that. What is that special entry? Useless fellow. Yeah? Whether you are doing it intentionally or unintentionally, you are
They don't take, they assume that they receive for themselves.
correct. You do it intentionally or unintentionally. You are like compensation for unauthorized use of goods. What is unauthorized use of goods? You give your bike for repair. Now the repair Anna will take your bike and use it as Rapido inside the city. Okay, ma. 5 people I'll bita can go. Okay, huh? You're happy, huh? No, no. That is what they're telling you. Unauthorized use of goods means I'm giving it to you for a specific purpose. You are not supposed to use it for some other purpose. To demand back the goods. Kulda. Right to accretion to the goods bailed. What is this? Again, exam question back. Again, one more brainy question. This cow and calf. Yes, Aduda. Now, people, what is it? Right to accretion to the goods bailed means people. I gave you one. That became two. You have to give me two also, not only one. Exam question. They gave a pregnant cow. There was a calf. You can't just give me back the cow when you can't keep the calf. You need to return both. Clear, huh? Hey, exam question, now people, next one. One more question that they can see is, imagine movable goods. Shares can also be considered as goods. Now, I was not in India, NRI. Yes, NRI gives shares to you to manage. Macha, you please take care until I come back. I gave you 100 shares of Infosys and I went. Now it's been 10 years. In 10 years, you tell how many times bonus issue would have happened. How many times dividends have been issued. Share split. So many things would have happened. Now when I come back, you're giving me back my 100 shares only. Is it fair? No, no. That is a right of accretion. Dividends are done. Bonus issues have been made. For all that, I have a right to recover. Hello. Done. Next one. Duties of bailey. Macha, in exam, remember one thing. Opposite is the other person. Hey, right to demand back the goods. What is the duty of the bailey? Right to give back the goods. That's his right. Right. I have a right to get back the accretion now. Anana. Yes, inconsistent use. Can I do rapido? No, no. So, hey, of course not. His right will be his duty. If it is a non-gratuitous bailment, it is my duty to make the payment. It will be his right to take the payment. Correct? No. Okay, see, to take reasonable care of goods. Take reasonable care of goods. Don't misuse it. Not to set up adverse title. I take goods from you. I sell it off to someone. Can I do it? No. Return of accretion, return of goods, not to mix the goods. If Bailey mixes it, possible. Not possible. Impossible. Clear? Hello. X gave horse to B when B locked it in stable. It went to a Hariharan. Okay. Rights of bailey. Rights of bailey. What is rights of bailey? What is rights of bailey? Opposite to duties of bailey. Hey Bhagwan. Kya hua? Okay. to deliver the goods to any of the joint bailers. If there are 2-3 bailers, I can give it to any one person in return. It is valid. I need not give it to only one person. If there are 3 owners, I can give it back to anyone. That's okay. Right to indemnity. If bailer has no title and bailee delivers them back to bailer, what is this? Let us imagine Nitish is a thief. Nitish took one bike from some parking lot. He went to a garage and he said, Anna, remodel this bike. That means what? Change the color, change the paint. Now, people, the actual owner filed the case on this garage person. Now, because of that, he suffered the loss. Who will bear the loss? They're telling Nitish has to compensate for the loss which has happened due to him. It can happen, na macha. You know, in Darshan's case, the murder case, accused number 19, you know who is accused number 19? Accused number 19 is a person who cleaned the vehicle. You know what is the vehicle in which the dead body was taken? The dead body was disposed. They took it to one place, garage. They got it cleaned. Whoever cleaned it is accused number 19. How will he know? But you are a culprit. Understood? So can this happen? Yes, so can people file? Yes, so yes, Papa sir, here at shampoo correct. Understood? Okay. Third one, claim compensation in case of faulty goods. Important. Remember, exam point of view. Bailee gets a right if bailer fails to disclose the fault known to him. Now, what is this, people? Zoom car, we take a car on rent. Now, in this car, brakes are not working. Now, we use it. Of course, there is an accident. Now, because of this, there is a faulty nature of goods. Now, am I entitled for compensation? Answer is yes. Now, sir, Zoomka says, sir, we did not know. It was a genuine mistake. We did not know. Whether you know it or not, if you have taken money, you have an obligation to give a right goods. In exam, this only they will ask. So whether you know it or not, if at all there is a bailment for money, then you are supposed to give a goods which is free from defects. Sir, what if it was free? I took the bike from my macha. If macha says, macha, I did not know that brake did not work. How does macha's bike, how will it be? Macha's bike generally. You put the brake in Koramangala, it will stop in Jayanagar. Our bus. Correct or macha? To stop in Jayanagar, you have to put in Koramangala. Now, people, you tell me. Now, Macha says, I did not know that, sorry, the brakes were not working. But believing in that, Nitish took the bike. Nitish was going in 180. Indian, he was about to take off. He tried applying the brake. Brake did not work. Now, Nitish can hold Macha liable. The question is Macha aware of it? Is Macha aware of it? That's what they're telling you. If bailment is for hire, bailee is liable even if he is not aware of it. Zoomer. Whereas if it is gratuitous, meaning free, Macha is liable only if the defect is known to him. So if he knew that the brakes are not working, yes, you are liable. If he can prove that I was not aware, then people, you are not liable. Clear? Hello? Remember, exam, they can ask you a question here. Next one, claim extraordinary expenses. What is extraordinary expenses? We took Zoom car. In between, there was a engine failure. Now, I was somewhere in between Chennai and Bangalore. Where do I go? There was nearby garage person who said, Rara. Now, we went. I had to spend money. Who will pay for it? They're telling you extraordinary expenses. For that, I am not liable. I am liable for ordinary expenses like toll charges, petrol charges. That I am liable. Extraordinary, I am not liable. Hello. Right to apply to court to decide the title of goods. Nitish, remember that one, the bike, stolen bike. Now he has given the stolen bike to garage to remodify it. Now the actual owner also came. Macha 1 is the thief. Macha 2 is the actual owner. Whom should the garage person give the bike to? Macha 1 or Macha 2? Now he will say, Ayo sir, I don't want any risk. I'll apply to the court. So there are two owners. You tell me whom to give, I'll give it to them. That is what is this. Right to apply to the court to decide the title of the goods. Clear? Next one. Duties of bailer. To receive back the goods after time and purpose. Correct? Service is done. Go and get back the goods. To indemnify any loss suffered. Correct? Duty to disclose faults in the goods bailed. Correct? Macha, brake not working. Pay necessary expenses. Agreed? Indemnify the bailee for premature termination. Correct? What was this, sir? TTA. I got it back. I said 2 years I will give. I got it back in 6 months. He washed and all that expense 40,000. Have a right to get it back. No, hello. Next one. Termination of bail. Right to lien. What is right to lien? Withholding the property which belongs to someone else until the payment is made. There are two types of lien. One is called as particular lien. One is called as general lien. What do you mean particular lien? Only when service of skill or labor is involved, right to retain until remuneration is received. Simple. I've given my bike for repair. I was not able to give back the repair charges. Now, if I do not give back the repair charges, he will not give me my bike back. Now, that is called as what? He has a right to lien. And that lien is called as particular lien. For that bike's charges, he can keep that bike until I make the payment. Whereas there is something called as general lien. What do you mean by general lien? General lien means nothing but people, bankers enjoy it. You know what do you mean by general lien? Let us imagine I have my FD with ICICI Bank. And from ICICI Bank, I've taken one more loan. Now, these are two different contracts. Agreed? I have FD, which I have opened long back. I've taken loan recently. It's a new contract. Now, I did not repay this loan. I did not repay this loan. Macha, bankers have a wonderful right. What is that called? Whatever is the loan I need to repay, I have not repaid. No, they can adjust one product to another product. They have my FD account, right? That FD account money they can take, they can set it off to this loan account. They have that right. If you have that right, the right that you have, that is called as what? General lien. Particular lien means what? For that product, you can only enforce and you can exercise your right only with that product, not with any other product. For example, to understand this, let us imagine Nitish has given a bike for service. Which bike?
KTM Duke.
KTM Duke. Now Nitish has one more scooty also. Which one? TVS 50. Yeah. Yamaha. I'll find ya. KTM Duke. Yamaha. Now there is one scooty, one bike. Correct? Huh? Now first what happened, people? First he gave KTM Duke. So he gave it today. He said, come back tomorrow. He went back. The bill was, people, 2,000 rupees. Now tomorrow he said, I want to give one more bike for service. That was Yamaha. So he took Duke and he gave Yamaha. And he said, I'll pay everything at once. Now, after 2 days, he again went. The total bill was, people, let us imagine, was around 3K. 2K for Duke, 1K for Yamaha. Now I went, people, when I asked the bill, he's saying 3K. I said, hey, 3K no, I'll not pay. Maximum I'll pay everything together is 2K. He said, if you don't pay, I will not give you your bike. He said, I'll give you 1K. That Duke you have charged more. I will not give you for that. He said, no, no, you have to give. He said, if you don't give, I'll not give your bike. Now, people, Nitish paid 1K, but Nitish is not okay to pay 2K for the Duke. Nitish is not okay to pay 2K for Duke. Now, what is the garage person saying? Until you pay the 2K, I will not give you this Yamaha bike. Are you okay? Are you okay? Can he do it? Remember, people, by default, not everyone has this right. What do you mean by particularly? The money belongs to Duke. You have a right to keep Duke only with you. You cannot keep Yamaha with you. That product's money should be kept for that product only. You do not have a right to cross change it like bank did. FD can be replaced with their loan agreement. But here, why can't he do it with Yamaha with Duke? Because Yamaha is there, he can hold it, no? That is the difference between particular lien and general lien. Particular means for that product, that money. General lien, any product, any money can be set off. If I have some other product belonging to you for some other contract, I can set it off. I have that right. Which you don't have it in the case of particular lien. General lien you can. Remember, by default, general lien will not be there with everyone. Only few people enjoy general lien. Who? Best example for you is bankers. If I have taken loan from them, I have my FD with them, savings bank account with them, my salary account is with them. They can take that money for the loan I need to repair. But Papa, our garage Anna, does not have that right. But if he wants to enjoy that right, he should specifically mention it in the contract that I will enjoy general lien, and we should have agreed. If you have agreed, yes, you enjoy. If not, you cannot enjoy. Understood? That's the difference between general lien and particular lien. And who else will enjoy this? Factors. Who is a factor? Factor is nothing but a business agent. Next one is war finger. What is war finger? Go down person. What do you mean by go down person? Let us imagine in go downs, it generally happens, no? In business. Imagine I have one goods. I would have kept it in one go down. Now, next month, that goods will be sold. I will replace it with another fresh goods. So, the goods are sold, but I have not paid his rent. The next batch of goods are kept. He's telling until you pay the previous money, I will not give you these goods. By default, the go down people have the right of general lien. So for the previous transaction, I can currently, whatever the goods I have, I can withhold those particular goods. Understood? Hello? War finger, attorney of high court. Attorney is what? Advocate. Meaning what? Let us imagine I get your court's judgment. So attorney is what? Lawyer. All this they will not ask. Okay. A is fighting his case in court. He cannot go directly. He is going through his lawyer. Now, A has not paid his fees to the lawyer. But lawyer has all the legal documents of this case. That is the court documents. You won the case. That verdict, judgment, all that is with B. They're telling you until he settles all your payment, you can keep all those documents belonging to A with you. It is allowed. That is the meaning of attorney of high court. Understood? Okay, next door. Policy brokers, again, nothing but insurance agents. If at all you have to pay some money to them, you got some insurance money. Whatever is the money you need to pay to them, they can withhold the money from the amount settled to you. They can withhold it. That is allowed. Alone are entitled for such lien. By express agreement, others may also have general lien. Garage Anna can have it, provided there has to be an agreement between the parties. Clear? Hello? Okay. Termination of bailment, how can it come? On expiry of the period stipulated, if I have given it for 1 year, 1 year is over, bailment comes to an end. on fulfillment of purpose. That means I've given it for repairs. Repairs is done, bailment comes to an end. By notice, gratuitous bailment people, anytime it can come to an end. I'll give you the notice, I can take it back. Non-gratuitous people, I cannot prematurely terminate it. The only ground when I can prematurely terminate it is inconsistent use. Correct? Zumo, Paramatma. By death of bailee or bailer, in case of gratuitous bailment, a person dies, the bailment comes to an end. On destruction of subject matter, Nitish gave his bike to Macha. Macha has parked the bike in front of his house. Earthquake came, earth split, bike went inside, earth came back. Destruction of subject matter. What will happen to the contract? Contract will come to an end. Void contract, no. Hello. Okay, the last contract in this is called as people pledge. What do you mean by pledge? Pledge is also a bailment only. Bailment for security is called as a pledge. For example, you want loan. You go to Muthoot and I give you gold. What will Muthoot do? Muthoot will give you a loan in return. Now, this is only called as what? You have given your gold to them. You have given your gold to them. Are they the owners? Are they the owners? The possession will be with them. If you do not pay the money, loan on time, then yes, they will sell the gold, they will recover the money. Now, people, this what you did is called as what? Pledge. Your gold is with them. That's why it's called bailment only. But why did you give it to them? It's for security purpose. That's the definition of bailment. Bailment meaning pledge is nothing but bailment of goods as security for repayment of debt. Hello? Essentials. Bailment for security, subject matter is always movable. Correct? Remember, land and all cannot come here. You can still take loan on land, but it will come under mortgage. Act only is different. It will not come here. Clear? Delivery of goods from pledger to pledgee. Bailer, bailee. Pledger, pledgee. Whatever are the rights and duties of bailer, bailee, write down same thing. It will be work same only. Nothing will change. If you guys are not able to remember. Hello. Okay. Pawnee's rights, that is nothing but pledgee's right. Right to retain pledged goods. Correct? So Muthoot, what are the rights of the Muthoot? Until you pay me principal, until you pay me the complete interest, until you pay the expenses on it, I have a right to keep the goods with me. If you do not give the money on time, I will not give you back the goods. Agreed? No? Right to retention of subsequent debt. What do you mean by right to retention of subsequent debt? Now, I have given you two debts, 1 lakh and 3 lakh. For this 1 lakh, I have given gold. They're telling you, I can keep this gold until you repay the second debt also. Something similar to general lien. The pledgee has the right, it seems. Until my subsequent debt is also repaid, I have a right to keep your goods with me. Hello? Right to extraordinary expenses. He can't retain the goods for it. What do you mean by the extraordinary expenses? Imagine to maintain this gold. If I incur any extraordinary cost, you cannot recover that cost from me. For example, safe keeping the gold is an ordinary cost. I can charge it for you. That comes under expenses. Polishing the gold is not an ordinary expense. It becomes an extraordinary expense. That I will pay for it. But if I don't pay for that extraordinary expenses, you cannot keep the gold with you. That will not have any right, but I have to repay. But if I don't repay, you cannot keep the gold for it. But ordinary expenses, until I pay the money, you have right to keep the gold. Extraordinary expenses, until I pay, you don't have right to keep the gold with you. Is this clear, all of you? Okay. Next one. When pawner makes default, what do I have a right? So if I do not repay the loan, I have a right to file a suit. Suit means file a case, and I can retain the goods with me only. Or I have a right to sell the goods after giving the notice. Meaning Muthoot will tell, sir, today is the last day. If you do not pay the loan on time, we are going to auction it. Now let us imagine the value of the loan was 1 lakh. I gave you the notice, you did not pay. We auctioned it. The gold, we were able to sell it for 80,000. First scenario. We were able to sell it for 1,20,000. Second scenario. Whenever there is a loss, I have a right to recover. Whenever there is a profit, I have to repay it to the pledger. Profit also I can't keep. Loss also I can't keep. I can only take what belongs to me. You take principal, you take interest. Anything extra, you have to repay it to the pawners. That is nothing but pledger. Understood? Hello? I hope this is clear. Okay, duties of pawner, liable to pay the debtor, of course. Disclose all the faults. If there is any defects in the product, you have to disclose. Pay extraordinary expenses. Indemnify pawnee if loss occurs. See, same thing only, no? Pay deficit if pawnee sells the goods, correct? No, see? You will pay, no? Hello? Okay, the last topic is pledge by non-owners. We'll do this along with Sale of Goods Act only. We have there also, no? Who can pledge it? Nemodat quad non habeta. Same thing. Again, the same topic only will come. We will do it when we are doing that. Yes, sir. Okay, let's last thing. Let us finish up. Agency. What do you mean by agent? Agent. Who is an agent? Whenever a person cannot directly act in lot of cases, what do? I appoint someone else to act on my behalf. Now this person is called as principal. This person is called as agent. Agent will act with the third parties. That is the outside world. Any contract entered between agent and the third party, any profit, principal only will take. Any deficit, also will be on the principal. Profit also on principal only. Deficit also on principal only. Agent has no liability. Agreed? But when will be agent liable? In some cases, the agent will be liable. When? Now, principal has clearly sold. I'm giving you my car. Can you please sell this car for a value not less than 5 lakh rupees? Agent sells it for 4 lakh rupees. I have clearly given you a scope, authority. And what you have done? You have sold it for a price lesser than the price I told you to sell. For the 1 lakh rupees, agent is liable. You have to repay that money to the principal from your pocket because there was a clear scope defined. In that case, agent will be liable. If not, principal only will be liable. Is this clear, all of you? Hello? Understood, Lila? Okay. So, agent is a party's principal, no? Agent. Can agent be a minor? Can agent be a minor? Can agent be a minor? Agent. Agent can be a minor. Okay. Can principal be a minor? No. Agent can be a minor. But remember, in our previous example, agent sold the car for 4 lakh. Technically, there was an obligation to sell it for 5 lakh. I sold it for a price lesser than that was told to me. The 1 lakh loss will be on the principal only. Agent will not bear it. If agent is a minor, there will be no liability. Agreed? This is what you saw under minor agreement. Agent can be a minor, but no personal liability. Hello? Okay. How is an agency created? First one is by express authority. This meaning a minor. No. See, by default, whatever the agent does, it is principal's liability. In that case, the agent is a minor. So minor has no liability at all. Yes, sir. People express authority. What if agent was insolvent? Meaning no, agent cannot be an insolvent person. Yes, sir. Now, express authority. On the spot, no, he cannot be. Yes, sir. Express authority. Now, how can we appoint an agent? One is express authority. This is only called as people power of attorney. I will sign from today whatever decisions taken by Mr. A, whatever he takes, I will be liable. Expressly, I'm saying, oral or in writing, it is called as express authority. Easiest way to appoint an agent. Second one is called as implied authority. What is implied authority? Based on circumstances. What is based on circumstances? Meaning nowhere I have clearly written, but the actions are such that on behalf of one person, the other person is always acting. So we will now estoppel will come into picture. Yesterday's mobile case, if you remember, when I started selling his phone, he did not speak. I will be deemed to act as an agent. He had a right to stop. He did not stop. Based upon the conduct, I become an implied authority. I become an agent. Third one, estoppel. Same. Hello. Fourth one, no. Necessity. What is necessity? Necessity. Correct, sir. Principal has appointed agent to do certain activities. But if at all there is any emergency, now agent can go beyond the scope. Whatever agent does, principal will be liable. Now, emergencies means what, people? Emergency means, remember, agent should not be in a position to communicate to the principal. And agent should have done whatever is the best alternative available. If I have done that, then yes, people, whatever actions agent did, principal is liable. For example, I tell you, there was a principal was sending some goods from one place to another place. Let us imagine from India to some other place, say Dubai. He was sending ship. In that, all those big containers are there. Hello? Agreed? Now what happened? We have appointed an agent to take care of this entire transaction. There is a, let us imagine a captain. Now what happened? In sea, there is a big tides coming. Now the ship, it became literally unsafe. I don't know if you guys know, it is a real life scenarios. Whenever the tides become unsafe, there will come scenarios that they will have to unload certain containers into the sea. They will have to push. They don't have a choice. Now, to save the entire container, now from there, which network will work? Geo will work. I'm not able to contact the principal. Now, whatever decision is taken by this captain of the ship, principal is liable, even though it can cause you a heavy damage, 50 crores you might lose. But at that point of time, that is the best alternative I could think. You are liable. That is only called as agency by necessity. I did not have power to push the goods into the sea, but now I got the power. Even though it is not there in my scope, I have it. I have the right to do it. Understood? Yes, sir. Next one, ratification. What do you mean by ratification? Now, for example, let us imagine there was Nitish and there was Macha. Nitish, okay, Noda? Now, Macha had one big building. Macha said, Nitish, I'm going for UK, NRI. Can you take care of my building? What did Nitish say? Hey, okay, Macha, Goda, I'll take care. Macha, nothing, the full building. Simply appoint one caretaker, let him just clean and maintain it. After 3 years, I'll come back. Nitish said, hey, Macha, Goda, I'll do it, not a problem. The moment Macha left, Nitish came and saw the building. Ayyo, in the prime center, this building, why to leave it idle? What did Nitish do? Nitish started a rental business there, meaning he started giving that property on rent. Let us imagine there are 3 floors. The total property is giving him a rent of per month is around 3 lakh rupees. So for 3 years, how much? Maths, better. For 3 years, let us take total is around 1 crore. That's the money you get. Yes, sir. Now, people, what happened? Now, Macha came back from UK. Now, he has come back. Now, people, the question is, Macha came back. Macha was expecting the building will be little beautiful. But whenever he came, what happened? In front of the building, one wire is there, full butter. That wire has become a smiley. Yeah, so much of clothes, so everything. Gate is so gate broken only. The people, Macha literally went, he was about to hit Nitish. Nitish took and gave one suitcase. Suitcase full of money. Now, what will Macha say? You only tell me. Macha will be angry or Macha will be happy? How much money? 1 crore rupees was given. Now, Macha will be happy or not? Yes, sir. Now, Macha has only one question. Now, Nitish, did you have this right to give this property on rent? You had the right. No. When you did this business, you did not have the power. 3 years is done. Everything is done. After Macha came back, Macha has a right. What? He can say yes or no for whatever has happened in 3 years. If he says yes, the entire 1 crore will go to Nitish. I mean, to Macha. Because I'm ratifying it. You did not have a right. Later, subsequently, I'm giving you a right to do all of that. Now, this is only called as what people? Ratification. Now, what if Macha says no? How dare you did it? Now, people, Nitish is right. You take everything. You make sure that the entire building is the same way when he left, however it looked. It is your duty to put that building in that place. Of course, Macha will definitely say no, he will take it. That means what? Along with that 1 crore, it is your duty to take the liability of the gate and whatever are the fixture mistakes, everything you have to bear it. It can come to 10 lakh, 15 lakh, you have to bear it. Agreed? This entire thing is called as ratification. Any doubt? Hello? Remember, for ratification, you should be aware of the complete knowledge of the facts. Hello? Now, for example, imagine in this ratification, the 2 floors gave him 40 lakhs, but the 3rd floor gave him 60 lakhs. Why? On top, Anna has done gardening. What gardening? Okay. Illegal law. Macha has done something illegal. Even though our Nitish has done it. Nitish has grown something because he got higher rent. He thought aesthetically it look good. Vastu. Now, people, even though Nitish has done it, Macha has no right to ratify it. You can never ratify an illegal act. Understood? Hello? Act should not be void or illegal. Clear? Hello? Okay, done. Ratification. Next one, appointment of sub-agent. Who is sub-agent? Delegators, non-potest delegate. Principal gives a duty to agent. Duty, the agent is a lazy fellow. He tells, I'll appoint one more assistant. He will do it. They're telling you people, remember, the generic rule is that delegators, non-potest delegate. What do you mean by that? A delegatee cannot further delegate. I've given on self some confidence, I'm given the work to you. You cannot further give it to anyone else. That right you do not have. Hello? But this rule has certain exceptions. What is that exception? So validity, generally you cannot do it. But what is the exception? Meaning, in these cases, even if you are appointing a sub-agent, it will be considered as valid. When people, if the terms of appointment allowed it. What do we mean by that? Clearly, while appointing the agent only is telling you, sir, I cannot handle it alone. I will appoint one more person. Are you okay with it? If he has agreed, people, then yes, you can go ahead. Next one, people, custom of trade provides for appointment. What is custom of trade provides for appointment? The business we are in, appointment of sub-agent is understood. Sir, how is that, sir? Now, a person is getting married. He goes and gives a contract to an event planner. Now, event planner, what he will only do? Cooking, anchoring, MC, dance, song, everything he will only do. No. It is understood. If you give it to him, he will further appoint the best chef. He will further appoint the best anchor. He is an agent. He is further appointing the right people for that particular task. If anything goes wrong, whose liability? It is his liability. The event planner's liability. It is event planner's liability. Now this is called as what? When the custom or trade allows it, it is understood. It is how it is. Appointment of sub-agent is valid. The third one, people, unforeseen emergency. We had given it to an agent. Agent is not able to do it. Let us imagine due to health issues. In that case, if he has given the work to someone else to get it done, it will be still valid if it is only in the case of emergency. Clear? Hello? Then third one is called as people substituted agent. What is the difference between sub-agent and substituted agent? Exam important. Substituted means what is substituted? Principal will come for agent. Sir, I want this work to be done. Agent will say, yo, sir, I don't know how to do it. Do one thing, you call him. So this person is called as substituted agent. What is the difference between sub-agent and substituted agent? In sub-agent, P has appointed A has appointed B is reporting to A is reporting to P. This is sub-agent. Substituted agent, P came to A referred B. Now B and P are doing the business together. They are directly related. There is privity of contract between them. They are directly related now. So this is called as what? Substituted agent. For whatever B does, P will be liable. Whereas here, for whatever B does, P is not liable. A is liable. Hello? That's the difference. Sir, in substituted agent, is A liable for anything done by B? Is he liable? Yes, sir. When, if at all, I referred a person without doing or without having due care, negligently I referred, or I referred for money. Why did I give B's contact? Because I will get some 10% commission. I did not give the best contact. I gave the contact which will give me commission. If I refer such people, then anything happens, I will be liable. A will be liable. If you do not refer a person in a good interest, negligently if you refer, you will be liable for whatever liabilities that happen in that contract. A will be liable. Are you getting the point? Hello? But if you have referred in a good interest people, A's liability will come to an end. Agreed? All of you? There is a privity of contract between B and A. Always remember. I mean B and P. Next one, right of an agent. What is the right? I have a right to get remuneration. Hello? Right to retain out of sum received on principal account. Advances made, expenses incurred, remuneration payable. What do you mean by this? Right to lien. If at all my remuneration is not paid, or if I have made any expenses from my pocket, if the principal does not pay for it, if I have your goods with me, I will keep the goods until the money is paid. There is nothing but right to lien. Hello? Next one, agent's lien on principal's property. Condition, lawfully entitled property should belong to the principal. Agent has particular lien. Right is lost. When possession is lost, agent waives his right or contract to contrary. Now what is that, sir? I have a right to lien, provided the product has to belong to the principal and I should be lawfully entitled to it. Now this right will come to an end if the agent has given back the goods to the principal, or this right will come to an end if the agent gives up his right. That time lien will come to an end. If not, agent will enjoy a particular lien, meaning I can keep the goods until the money is paid. Clear? Okay. Next one, sir. Right to indemnity. For lawful acts done in good faith, non-liability of employer of agent to do criminal act, Compensation for injury caused by principal's neglect. Now, what do you mean by that, people? Imagine principal gave an agent to sell a car to third party. Now, whose car was this? Principal had stolen it and I gave it to an agent. Agent sold it to someone. Now, he filed a case on agent. Agent will not be liable. It is a right of the principal. I mean, it is right of the agent to get indemnified. If someone files a case on me for acting on your behalf, if I suffer any loss, it is your duty to make good the loss. You have to pay for it. Agreed? Yes, sir. And no, and remember one thing. If at all there is employer-employee, if there is an employer, there is employee. If employee does any criminal act, what do you mean by that? Imagine if this person does any murder. For that, employer will not be liable because generally what did we say? Principal agent. If agent does any criminal act, principal will not be liable for the criminal act. It will be the agent's liability. You will be arrested and not the principal. That's what they're telling you here. Non-liability of the employer of the agent to do any criminal act. Whose liability will it be? Who will be arrested? It will be the agent who will be arrested. Criminal act, it's your act only. Clear? Hello? Compensation for injury caused by principal's neglect. Same thing. Now, imagine I told principal said agent, you go and get some contracts from the retailers. I will supply you some goods. Now, agent went and entered into a contract with retailers, but principal did not supply the goods. It is your neglect and agent suffered the loss. It is my duty to pay for the loss suffered by the agent. Whatever we saw in the previous example, same thing. Next one, duties of agent. Duty to execute mandate. What do you mean by duty to execute mandate? Principal clearly told, for whatever the goods we have in go down, take insurance on it. It is your duty to take insurance on it. If you don't take it, any loss happens, agent's liability, it will be. Remember, exam question. Principal told an agent to insure the goods they have. Agent failed to take an insurance policy. The next day, the goods were damaged. It was considered the entire damage will be borne by the agent and not by the principal. Clear? Next one, duty of reasonable care and skill. What is the duty of reasonable care and skill? Meaning, people, principal told agent that can I make a credit sale? Meaning, cash sale, credit sale. You can make a credit sale. Principal has given you a right. But that credit sale when you're making without taking cash, if you're giving credit to someone, it is your duty to take reasonable care. You have to know the background of the buyer. You cannot give credit period for everyone. You can only give it to those people whom you know, whose credit worthiness you know. If you give someone credit just because I allow you to give, if something happens, then agent will be liable. That's the meaning of it. It is your duty to take reasonable care. Hello? Sir, what if the principal has not said anything that I can give the goods on credit or not? Then in such case, what to do? You follow your instructions. If instructions are not there, follow customs. Custom means what, people? You follow your industry. You go to hotel. Will you get food on credit? Answer is no. That's the custom of hotel. You do not have it. So follow what your industry follows. Clear? Okay. Compensate principal if acted otherwise. So agent, if he does not follow it this way, it will be agent's liability. Next one, avoid conflict of interest. What is this? Principal told agent to sell my car for a good price. Now, what did agent do? Agent sold the car to the third party. To whom did he sell? He said, give it to me in a reasonable price. I'll give you 10% as commission. Principal gave his car to A to sell it. Agent is selling to a person, whoever is giving him good commission. That is what is called as, people, avoid conflict of interest. That is nothing but we had already seen also. What is that? Interest against obligation, opposed to public policy. You're not supposed to do that. You're supposed to do what is beneficial to your principal and not what is beneficial to your pocket. Hello? Next one, communicate with principal in difficulties. If you're not able to make decision, call and then take a decision. Not to make secret profits. See, if this is there, intimate and do. Don't do it without intimating. Next one, to render proper accounts, have a proper accounts. Whenever asked, give it. Not to delegate, whatever we saw. Generally, principal will appoint agent. Agent cannot appoint a sub-agent. This is a general rule. But of course, there are exceptions which we saw. Pay sum received for principal. If I have received anything in the business, it is my duty to give it back to the principal. Not to use confidential information against the principal. So, if for example, you are CA, you will be getting all your clients' data. Can you go and give it to the competitor? That's what they're telling you. You're not supposed to do. Next one, principal or agent's liability to third parties. Who are liable to principal or agent? Principal or agent? Generally, people, it is principal's liability if agent is acting within scope. If agent is acting beyond the scope, who will be liable? Agent will be liable as long as agent is not a minor. Agreed? Agent is not personally liable, but for this there are exceptions. What is that? This can be an example. I mean, this can be, you can expect a question here. Generally, it is principal's liability. But when will it be agent's liability? Whenever you are a pretended agent. What do you mean pretended agent? The world does not know that I am an agent. Now, for example, in this case, people do not know that he is the owner. They thought I am the owner. Now, if any loss happens, they will come and file a case on me and not on the principal. That is the meaning of pretended agent. Are you getting the point? Hello. Foreign principal. What is that? Principal stays in foreign country. Agent stays in India. Anything happens, where will I go and file a case on the principal who is outside India? I will file a case on the agent who is in India. In this case, agent will be liable. Third one, agent does not disclose the name of the principal. Meaning, there is a principal, there is a agent. Agent is never disclosing the name of the principal. If you do not disclose who is the principal, then agent only will be liable. Whom else I can file a case on? Next one, incompetent principal. Minor, we have already seen. If any act is done by them, then they will always be, agent will be liable. It will not be technically minor also. This example can be a person who has become insolvent. If a principal becomes insolvent or a principal becomes unsound mind, who will be liable? Agent will be liable. Correct? Next one, principal's liability when agent exceeds authority, which we have already seen. If agent exceeds, what will happen? So it depends. Let us imagine if agent, I told agent to buy 1000 kgs of raw material. Agent has purchased 1200 kgs. This contract can be separated. No, up to 1000 kgs, principal is liable. 200 kgs, agent is liable. I told my agent to buy a car for 5 lakh. Agent has purchased the car for 10 lakh. Can I separate it? First 2 wheels you use, next 2 wheels I use. Can I separate it? No. When the contract cannot be separated, the liability of the entire contract will be on the agent only. That is what is written here. If it is separable, principal will be liable to the extent authorized. Non-separable, agent will be personally liable for the entire contract. Car example. Hello? Any notice given to agent is equivalent to giving it to the principal. If third party wants to communicate anything with the principal, communicating with the agent is like communicating with the principal. Effect of misrepresentation or fraud by agent. What do you mean by this, people? Principal gave a car to the agent to sell it to third parties. Now agent sold it. How did he sell it? The mileage of a car, people, it is coming to say, for example, 12 kilometers. But agent, for the purpose of commission, he said, so the car gives you 25 kilometers mileage. Now agent has done fraud. Let us imagine there is no way that the buyer can make it out. There is a defect in the meter or something. He cannot make it out. The question is, who is liable for this? Agent is liable or principal is liable? For whatever the fraud done by agent, who will be liable here? Principal or agent? Principal or agent? Remember people, it is my duty to appoint a proper agent for any word he uses to sell this car. The liability is on me. It is my duty to appoint a right person. Who will be liable? Principal will be liable. Why? Because it is within the scope. I told him to sell the car. He is selling the car. Hello? So whatever I have authorized him to do, if he is doing, and if he uses any fraud, misrepresentation there, the liability will be on the principal, provided if it is within the scope. If it is beyond the scope, something which I have not authorized him to do, he is doing that. For that, I am not liable. But here, the buying of a car, I have authorized him. If he does something, I am liable. Selling the car, I have authorized him. I am liable. Hello? Understood? Huh? Next one, beyond the scope. Okay, that is what we have seen. Next one's the right of third parties. Contract made by a undisclosed agent. If agent does not disclose that he is an agent, if principal is disclosed before contract is completed, the third party may refuse to fulfill the contract. Now, what do you mean by this? If agent does not disclose that he is an agent, if principal is disclosed, now what do you mean by that, people? Let us imagine there is a person. He sends his agent to the bank to get a loan. Now, people, the banks, of course, whenever someone is coming for a loan, the banks will be happy. The banks will say, sir, please come and sit. They'll give you the loan. Yes, sir. Everything is okay. Now, who is he? They are only contacting with the agent. They have not yet seen the principal. At the last day, people, the agent will tell, sir, you know for whom I'm taking the loan. They asked for whom. Sir, we are taking the loan for Vijay Mallya. Now, people, if at all the third party gets to know the principal's name after entering into a contract, the third party has a right to cancel the contract. They can rescind it. That's what is written here. Read. If agent does not disclose that he is an agent of Vijay Mallya before the contract is completed, the third party may refuse to fulfill the contract. I can say I will put an into this particular contract if I get to know who the principal is. Hello? The third party has this right. Next one, what else right I have? Right of third party. Performance of contract where agent is supposed to be principal. What do you mean by those people? Agent, in my case, I told you this, estoppel. Agent is assumed. People do not know that principal even exists. People are thinking principal, I mean, the agent itself is the owner. In that case, people, the third party will file a case on the agent only. If I need anything, I will come and ask the agent only because I don't know who the principal is. Because the world is assuming that the agent itself is the principal. That is what is this? Performance of contract where agent is supposed, meaning assumed to be the principal. I will come and file a case on the agent only because I don't know who the principal is. Hello? Next one, option of third person to sue the agent or principal. So the third party has a right. In some scenario systems, I can file a case on either agent or I can either file a case on principal. It is my choice. When will I get this right? First one, cases where agent is personally liable. Where was the scenario where agent was personally liable? These scenarios. Now it is a third party's choice. If they want, they can file a case on agent. If they want, they can file a case on principal. It is their choice. When else they can file a case, whether on agent or principal? Consequence of an inducing agent or principal to act on a belief that principal or agent will be exclusively liable. What do you mean by that? Sir, there is a principal who has given his car to the agent to sell it to a third party. Now we all know that this car does not belong to the agent. But the agent has clearly told, sir, you take the car, you use it. If you have any problem, you come to me. Agent has given you a belief that anything happens, you come to the agent. If they have given you that belief, you will go to the agent only and not to the principal. So when an agent has given you, induced you, saying that if there is anything, you come to me, he will come to you only, not to the principal. That's the meaning of what people, consequence of an inducing agent to act on the belief that agent will be exclusively liable. He said, you come to me, I'll come to him only. Or if principal says, you come to me, I'll come to him. That is what they're trying to tell you. In certain cases, a third party will have a option whether to go with principal or the agent. These are the scenarios. They can ask you a question here. Remember and go. Clear? Hello, hello. The last one, termination of agency. When will the agency come to an end? First one on completion of business. I told you to sell the car, you sold the car, agency will come to an end. Next one, expiry of time. I appointed you for 1 year, 1 year is done, agency will come to an end. The third one, principal becomes insolvent. Of course, agent will be liable for that contract, but the contract after that will come to an end. Contract will not continue beyond that point. Next one, revocation by principal or renunciation by agent. Revocation means what? I appointed you for 1 year, but in 6 months only I'm taking back my right. Principal is taking back the agency. That is the right I've given you, I'm taking back. When principal can take back, agent also has the right to give it back. So this is like people removing. This is people like resignation. That is only called as renunciation by agent. You have appointed him, but he is giving up the right. Next one is death or insanity of principal or agent. Whoever dies people, the agency will come to an end. But remember, whenever there is revocation or renunciation, meaning you were appointed for 1 year, you are taking back in 6 months or he is giving back in 6 months, it will be considered as breach of contract. If there is any damages, you are liable to pay because you are giving up in between. That liability will always be there. Hello, correct? But when will this revocation be effective? Meaning, I have appointed the principal has appointed the agent for 1 year. He has appointed the agent for 1 year. Now, I communicated in between that I am taking back the agency. When did I communicate? I communicated on 1st May 2026. Hello? Now, I have communicated this to the agent. But agent has still acted on behalf of the principal. He has acted till 30th May. Now, my question is, I have communicated to the agent on 1st May 2026 that the agency will come to an end. But he has still continued to act as an agent with certain third parties. Let us imagine there was a person called A. Okay, let us imagine we have entered into a contract with a person called B on 30th May 2026. For this contract entered on 30th May 2026, who is liable? Is principal liable or agent liable? Principal or agent? Principal has taken back the agency on 1st May. Contract was ended on 30th May. Very good, sir. Remember, people, for this contract, principal will be liable. Why? Your agency will continue until the third parties are also informed that the agency has been terminated. You have informed on 1st May only to the agent. Have you informed it to the third parties? If third parties are not aware, then you are liable as a principal until they are aware. So in this case, third parties were not aware, or are they aware? If they were aware, your liability will come to an end. If third parties were not aware that you have taken back the agency, then principal will be liable for the contract entered on 30th May. Exam, they can ask you, remember and go. Hello? Clear? Hello? Okay, go for a break and come. How much time? 1.5 hour. Why? Go 3 hours. Hey, 1.5 hour, that only will, you guys said you will sit for some time. 1.5 hour will be like what? 3 o'clock.
Sir, you have to go there and come.
Para. Hey, 1.5 hour is too much, da. Hey, 1 hour is also too much, da. Effect of termination of Madiko. When will it be effective? Agency comes to an end. Till 45 minutes. I 1 hour. 1 hour 15. Hey, it will be too long, da. 1:30, 2:30 it will go to. Okay, Madi. 2:30, I don't know the practical difficulty, but that's why I don't know. You're saying you have to go to, how many of them have to go to PG and come? Oh, then whole green, what else I can say? 1 hour 15 minutes, Okay. 2:30. Yeah, let's see some 2-3 more questions and then let's go for the next topic. Concentrate. Mr. Rich aspired to get a self-portrait made by an artist. He went to the workshop of Mr. C, an artist, and asked whether he could sketch the former's portrait on oil painting canvas. Mr. C agreed to the offer and asked for 50,000 as a full advance payment for the above creative work. Mr. C clarified that painting shall be completed in 10 sittings and shall take 3 months. On reaching the workshop for the 6th sitting, Mr. Rich was informed that Mr. C had become paralyzed and would not be able to paint for the near future. Mr. C had a son, Mr. K, who was still pursuing his studies and had not taken up his father's profession yet. Discussed in light of Indian Contract Act, can Mr. Rich ask Mr. K to complete the artistic work? Could Mr. Rich ask Mr. K for a refund of the money paid in advance to his father? Possible, not possible? Whatever advance was paid is supposed to be returned. That is liable. And is K personally liable to fulfill the contract? Answer is no, because it involves skill and confidence. The person himself has to perform, not legal representatives. Agreed? Mr. Murari owes a payment of 3 bills to Mr. Girdhari as on 31st March 2022. That is 12,120, which was due in May, 5650 August 2020, 9680 in May 2021. Mr. Murari made payment on 1st April 2022 as below without any notice of how to appropriate them. A check of 9680 was given, a check of 15,000 was given. Advice under provision of Indian Contract Act 1872. 3 loans were taken. He repaid these 2 amounts on 1st April 2020. How would you appropriate it? First one is for May 2021. If nothing is communicated, you will take it towards the third one only? Yes? The first one is for first one if nothing is communicated. Today only we did this example. Again, that only you guys will okay, see here. Hey, I told you whenever 4 scenarios, keep it in mind. First, the debtor will have a choice. Whenever debtor is silent, the next one check if circumstances will prevail. Circumstance means what? I'm exactly repaying 9680. There is exactly 9680 debtor. When circumstances show if everything is silent, then as per circumstance, you have to take it towards the transaction which is similar to that. We saw today only example, 35,000 or something was the example I told you. So 9680 will be taken towards the third transaction. If the debtor was silent, 15,000 will be towards what? First will be towards first transaction. Excess, if any, will be towards second transaction. If everything is silent, that is how you will take. If everything is silent, what will we do? The next option will be given to the creditor. The creditor can take in his choice. If creditor is also silent, then you will take it in FIFO method. But in this case, which one will creditor choose? Which one will he choose? It will definitely be which one? It will be towards first one only, because they are trying to ask you time bar data. 2018 it was taken now. You are in 2022. It's more than 3 years. So can you still take towards that? Answer is yes. So if creditor is given a choice, he will take towards the first transaction only. Hello? Had nice lunch, Pillow kodana? Pillow? Sir, that's the best. Hey, same question asked second time you're answering wrong means what do I tell? Okay, see. X, Y, and Z jointly borrow 90,000 from L. Decide each of the following in the light of the Indian Contract Act. Whether L can compel only Y to pay the entire loan of 90,000. Possible, Whether L can compel only the legal representatives of Y to pay the loan of 90,000 if X, Y, and Z died. Oh. If X, Y, and Z died, can they compel only the legal representative of Y? So all the legal representatives are liable, not only one legal representative. Agreed? Okay. Whether Y and Z are released from their liability to L and X is released from his liability to Y and Z for contribution. If L releases X from his liability and sues Y and Z for payment. Whether Y and Z are released from their liability to L and X is released from his liability to Y and Z for contribution. If L releases X from his liability and sues Y and Z for payment. Remember, if I release one party, you are liable for the other promisors. For the creditor, you are not liable, but for the other joint promisors, you are liable. You will not be relieved from the liability within you guys. The creditor may relieve you, but amongst you, you are liable. Meaning, if imagine if L is relieving X, Y and Z will pay his money, but Y and Z can recover that money from X, no? Correct. L, lender can say that you don't pay it to me, I will collect it from them. But amongst them, they will be liable. See, whether Y and Z are released from their liability to L and X is released from his liability to Y and Z for contribution. If L releases X from his liability and sues Y and Z, same thing only they are telling you. L is releasing who? X from his liability. Is he free from his liability to Y and Z? If I am relieving X, is he relieved from his liability to Y and Z is what they are asking. That only they are asking 3 times, that's all. Read, whether Y and Z are released from their liability to L and X is released from his liability to Y and Z for contribution if L is releasing X from his liability. Example, correct? I hope you guys understood. What they're asking you is simple. L is releasing X. Based on this, 2 questions they're asking you. Because of this, are Y and Z are also released? No, that is the first question. Whether Y and Z are released. Are they released? Illa. Okay, next one. And X is released from his liability to Y and Z. Because I released you, is X's liability to Y and Z? Is this liability released? That is what is the question now. What tricky? Understood? Yes, nice, no? Like this, you should solve. Okay. Mr. X and Mr. Y entered into a contract on 1st August 2018 by which Mr. X had to supply 50 tons of sugar to Mr. Y at a certain price, strictly within a period of 10 days of the contract. Mr. Y also paid an amount of 50,000 towards advance as per the terms of the above contract. The mode of transportation available between their places is roadway only. A severe flood came on 2nd August 2018 and the only road connecting their places was damaged and could not be repaired within 15 days. Mr. X offered to supply sugar on 20th August 2018, for which Mr. Y did not agree. On 1st September 2018, Mr. X claimed compensation of 10,000 from Mr. Y for refusing to accept the supply of sugar, which was not within the purview of the contract. On the other hand, Mr. Y claimed for refund of 50,000, which he had paid as an advance in terms of the contract. Analyze the above situation in terms of the provision of Indian Contract Act and decide on Y's contention. Read once again, of course. Understood? What is the answer? Supervening impossibility. Okay, I think they have asked more questions here. What and all? That's all. Supervening impossibility is the answer. Time is also essential. Okay, tell me the answer. Conclusion only tell me.
Why can claim the refund?
Why can claim the refund? Why can claim the advance amount back? Okay. X cannot compel Y to accept the goods. Void agreement. Void contract. That's the answer. Most of the think that's the answer. Hello. Mr. Y is entitled to the advance amount, but Mr. X cannot be entitled to compensation. The contract becomes void. Impossible to perform, so it becomes void. So can you show the answer? Okay. I'll share it with you. If you have not yet received it, probably wait till tomorrow. I'll add a few more questions and I'll share it together. I've added only till certain point. I think I'll send it at once. I'll send it at once. Yes, sir. Is the contention of Y correct? What is the question? And decide on Y's contention. What is Y's contention? Y claimed refund of 15,000, which he had paid as an advance. Can he get it back? Answer is yes, sir. Now look for your provision. What does it say? Impossible after entering into a contract. Can I say it as supervening impossibility? Answer is yes. Because of that, the contract becomes void. Because of that, there's a clear rule. Remember, if a contract becomes void, you have to write this point. Any advances, any money received, the person is supposed to repay that money back. Now, those grounds are to be mentioned. If you mention that, people, yes, sir, based on that ground, Y can be entitled for the refund of money allowed. Is this clear? If you write that entire thing, that is when you will get the mark. Supervening impossibility is one part. But on what ground is Y getting the money back? In void contract, it is written. If the contract is void, you get a right to take back the money. Whatever is given as advance. You answer the same thing in that painting case also, no? Until that point is written, you will not get that full mark. That is where they will deduct that 1 mark or 2 mark and all. Clear? Okay, A, B, C, and D are the 4 partners in a firm. They jointly promised to pay 6 lakh to F. B and C has become insolvent. B was unable to pay any amount and C could pay only 50,000. A is compelled to pay the whole amount to F. Decide the extent to which A can recover the amount from D with reference to the provision of Indian Contract Act 1872. Joint promisors. 4 partners together have taken 6 lakh. B and C has become insolvent. So 2 partners have become insolvent. B was unable to pay any amount, but C could pay around 50,000 rupees, it seems. A is compelled to pay the whole amount. So A only has paid 6 lakh. And what are they asking you? How much? Decide the extent to which A can recover the amount from D. What is the money A can recover from D is what they're asking you. Understood the question, huh? Joint promisors, one person was compelled to pay, he can recover the money from other partners. Now they are asking you what is the maximum he can recover. How much? They are asking you money. 2 lakh? Okay, 2 lakh 45,000. 35. 25,000. Okay. Huh? 1 lakh 25,000. Okay. Up to? No, there is an amount involved. Huh? 2 lakh 75,000. Whatever is the question, you guys answer for that. How much? How much? 2 lakh 75,000. 1 lakh 55,000. Sabash. That's how the competition should be. 2 lakh 75. 2 lakh 75. See, 2 lakh 75. What is that they're telling you people? See, by default, A's liability, everyone's liability is 1.5 lakh. Huh? Correct? Huh? Write it like this only and say, there is all the liabilities. Now, in that, one partner, we could not recover anything. From one partner, we recovered 50,000. That means what? His 1.5 lakh and his 1 lakh has to be shared between A and D. Agreed? Huh? That means what? 2.5 lakh is the money. Huh? Now 2.5 lakh divided between 2. How much? 1 lakh 25,000. Now D add 1 lakh 25,000 to D. 2 lakh 75,000 is what is D's share. Now what they have asked you clearly in the exam. What is the money I can recover from D? The money I can recover from D is 2 lakh 75,000. This is how you need to write. Yes, sir. Hello. See, same usual question, but the way it is questioned is different. That's why it was a good question. Okay. Correct? Huh? Okay. X entered into a contract with Y to supply him 1,000 water bottles at 5 rupees per water bottle to be delivered at a specified time. Thereafter, X contracts with Z for the purchase of 1,000 water bottles at 4.50 per water bottle. And at the same time, told Z that he did so for the purpose of performing his contract entered into with Y. Z failed to perform his contract in due course, and the market price of each water bottle on that day was 5.25 per water bottle. Consequently, X could not procure any water bottles and Y resigned the contract. Calculate the amount of damages which X could claim from Z in the circumstance. What would be your answer if Z had not informed about Y's contract? Explain with reference to the provisions of Indian Contract Act 1872. Huh? Huh? Up to 2,500. Huh? That's the answer. Huh? Any other answer? Total. Give me total. What is the maximum I can recover? Total is 2,500. Huh? Total is 2,500. Okay. 750 rupees. Okay. No, I'm asking. It can be right also. I'm just asking. Da. Huh? 5,000. Okay. 1,250. Very good. 1,250. Okay. 750. Okay. And 1,500. Very good. One question. 8 answers. Innu you guys will give me more. 750. Okay. Tell me first of all, on what basis? How much is the compensation you're claiming? Well, first of all, what type of damages? I hope all of us know it's a damages, breach of contract. What type of damage? Ordinary damage or special damage? Okay, first question is what? There are two questions involved. I hope you guys saw it. Don't tell me you saw only one question. There are two questions, Noda. Calculate the amount of damages which X could claim from Z in the circumstance. That's the first question. Second question is, what would be your answer if Z had not informed about the Y's contract? That's the second question. First question is special damage. Second question is ordinary damage. Whenever I've informed my purpose, then what I can claim from you? Special damages. The purpose is communicated. In the second case, because the purpose is not communicated, I cannot claim for that particular damage. So what I can claim is ordinary damage. Hello. What is the answer? The problem in the instant case, exam performing there is a knowledge of special circumstance. Hence, X is entitled to claim 500 at the rate of 0.5 paise. That is for 1,000 water bottles. Difference between the procuring price of water bottle and contracted selling price. Agreed, being the amount of profit X would have made by the performance of his contract. If X had not informed Z of Y's contract, the amount of damage would have been the difference between contract price and the market price. That is nothing but 0.75 paise, 750. And I don't know what you guys answered for. 750, if it is for this one only, okay. And I don't know where this 2,500, 5,000 and all came from. Yeah, but okay. You guys added it up. Oh, that's how you added and gave. You multiplied. Okay, ಏನೋ ಒಂದು ಮಾಡಿದ್ರಿ, but you guys understood, hello. Okay, we'll see this again later. We'll first go back there and we'll finish it off. Taka. People, yeah, people. Hey, people. ಯಾಕೋ ನೀವು they remembered easiest way to score more in law is open questions. Solve as many questions as possible. That's the easiest way. If you ask me shortcut, that's the shortcut. At least by the time you guys go to your exam, you should have at least written and solved from today. Take 3 questions a day. If that will take you to 100 questions in writing, do it. And when you're at least seeing questions and solve at least 200, 300 questions. Meaning I'm seeing, go through it the way we are doing it now. That's when you will be able to understand how to see that particular topic. The way you have understood versus in reality, what it is, you will be able to get the difference. Are you guys understanding? Hello? Okay. Because there's a lot of gap between what the topic is and the way you guys are thinking. I don't want to scare you and all. 1 month is there. Law, you are still thinking and struggling in fundamental questions. Good mindset, I don't know. But okay. Sale of Goods Act 1930. But I hope all of you are aware of the topics, based upon the reflection I get. I am feeling conceptually you guys are not up to the mark. Upfront, I'm telling you. Because my usual marathon is 11 hours. By today, we complete 11 hours. You're understanding something? That's what I'm saying. 11 hours are completed, but not the 11 hours was the topic. Yeah. I don't know. With most of you, I'm feeling that you're not aware of the concepts. With most of you, I'm feeling that. Even just now in the break, they were asking me, how is it? I said, no, it's not up to the mark. Marathons has to go like this. I'm explaining the concepts. Because when I say, you say, okay, you reply, you go, we go ahead. But you guys are even struggling at that point of time. Not scaring you, but don't go with that attitude. Because exam will be predictable, not surprise. Result should never be predictable. It should be a surprise. Correct? No. Attitude matters. In exam, result will not just like that come off. Especially, macha, once if at all you have gone and come back, then I'm saying you should wake up. I don't know how many of you have gone, you have come back, I don't know. But I'm telling you, wake up. Failing is not a problem. Failing in the same way again is a problem. You know what I'm saying? I know that if I go in this way, it's a dead end. Again, I'll go and see if the road is open means it's a dead end. If the road they'll open now. Yes. For example, you know today's marathon. You guys go home and try to read and come? No. Impossible. That's the difference between the previous batch and your batch. Meaning, if you read and come, the way you understand the concept will be different. That's not happening. Okay. After marathon, are you going and reading this only? Reading. From yesterday's topic only, I asked questions today. That only we are going wrong. Second thing I'm seeing is involvement is not there. What is involvement? I am doing, you guys are doing. You should be into the class. Don't take it as a formality. Yes. See, I'm not telling you, people, another one day, if I close my eyes, my batch is done. My burden is done. Not yours, no? Yes. You guys only tell. You don't tell it for me. Are you guys happy the way you guys are? Then okay, I don't mind. I'll be asking 100 topics. I'm telling this. I'm asking that. You guys will neither say yes nor no. An exam, 1 month. Yeah. I'm telling you people, miracles can happen in all other subjects, but not law. Trust me, miracle word does not exist in law. Unfortunately, it is built like that. Your yes or no conclusion will not give you a mark unless your provision is right. Second one, your writing matters. And yesterday only I told you, it will test your concept and language. We have to frame that also. How will you frame? Yes. Wake up, be a little more, probably a little more dedicated. Yes, as I always say, exam should always be a suspense, surprise. It should not be predictable result. Agreed? Okay, nonetheless. Okay, next one, let us start. Sale of Goods Act, formation of contract of sale. So goods, what is the definition of goods? Goods means all movable properties. It includes stock, shares, growing crops, grass, and things attached to the land agreed to be severed. Correct? It does not include actionable claims and money in circulation. That's the goods definition. It means movable property other than actionable claims because it is governed under Negotiable Instrument Acts. Actionable claim is nothing but a document which gives you a right to demand money from the other party, like promissory note, bill of exchange. Based on this, I can demand money from the other party. Next one is money in circulation. What is money in circulation? The currency which is existing and legal today cannot be considered as goods. What about currency which is not in existence today? Can be considered as goods. Example, antique coins. It's money only, but today it is not in circulation. It can be sold as a goods. Sir, and also includes stock and shares, growing crops, grass, and things attached to land. This is what I was telling you. Shares is considered as goods. Your shares, equity shares, is considered as goods. This was the first law that was applicable for share transfers. SEBI and all was not there, no. Where was SEBI? Where was SEBI in 1880? But still shares were there. 1920, 1930. Where was SEBI? 1992 SEBI came. 1956, the first securities related law came. 1956. Then until then, if a person wants to buy, sell shares and all, which law was applicable? Sale of Goods Act was applicable. Now we do not follow because there are more specific laws today. Yes, sir. Okay, growing crops, vegetables, grass, all things will come there. Next one, things attached to land and agreed to be severed. What is this things attached to land? Can I say trees attached to land? Is tree a movable property or immovable property? It depends on this. Agreed to be severed means what? There is sandalwood. A sandalwood is there. This person comes. It becomes movable property. Until this person comes, it is a immovable property. Agreed? Agreed to be severed means there is an agreement made to cut it. Until it is not cut or until there is no agreement, it is coming under immovable property. It will come under immovable property. The moment agreement is made, it comes under movable property. Best example is timber. What do you mean by timber? Timber means people, tree which is specifically grown for the purpose of furniture, construction. It is grown only to cut. They are considered as what? Timber. So once it is grown, an agreement is made to cut it. It is called as what? Movable goods. When it is called as goods. Clear? Hello? Okay, further classification of goods. Goods can be further classified into existing goods, future goods, contingent goods. Now, existing goods means what, people? The goods which are existing. Remember, how do we have to write it, people? The goods which are owned or possessed at the time of contract of sale is called as existing goods. Meaning what? When the sale is happening, people, the goods have to exist. When the sale is happening, the contract, that whenever you are entering into a contract, the sale is made. At that time, goods should be existing. It is already present. Such type of goods are called as existing goods. Existing goods can be further classified into three things. One is called as specific goods, unascertained goods, and ascertained goods. Now, what do you mean by specific goods? Which are identified at the time of contract of sale. Now, what do I mean by this? Now, whenever I go to a shop, a physical shop, I ask him, say for example, there is a lot of chips packets there. I go, I tear a chips packet I want, and I say I want this one only. Imagine there are so many flavors. I take the chips, which is say for example, green color. I'll tear it. There are so many green color also. I'll take that one which has full air. I'll tear it and I'll say I want this only. So when a contract is being made, I know exactly which chips packet I'm going to get. It is identified. When the contract is being made, you already know which product you are going to get. It's called as specific goods. So what if I ask for a chips packet, but the chips are behind the shopkeeper? There are some 50 packets behind the shopkeeper. Now you say, sir, I want chips packet, 10 rupees wala. Can you give me? He says, yes. Contract is made. Offer plus acceptance is done. But do you know which packet you are going to get? He goes inside. There are 50 packets. In that, randomly he tears one. He comes and gives it to you. Goods which are identified after the contract of sale is made is called as what? Ascertained goods. Sir, before the what is that packet was torn, it was there in that 50 packets were together in the bulk. The contract of sale is made, but the goods are not yet identified. It is still in the bulk. What do we call these goods as? Unascertained goods. The goods in the bulk which are not yet identified. They are called as what? Unascertained goods. After the contract of sale is made, if the goods are separated from the bulk, we call it as ascertained goods. Yes, one question you can expect. And remember, people will write the examples here. Remember, try to remember the definition. Unascertained, ascertained means what? The goods identified after the contract of sale. You have to write it like that. People will write something which is separated from the bulk. That is not a definition. That is an example. Remember and go. Okay, next one is called as future goods. What is future goods? Goods which are acquired, manufactured, produced after the contract of sale is made. A company called as Kisan Company goes to farmer and say, we want to buy tomatoes. Farmer says, okay, come back after 6 months. We enter into a contract today, but the crop will be produced after 6 months. Such type of goods are called as what? Future goods. Dana. Third one is called as contingent goods. What do you mean by contingent goods? Now, for example, there are these paintings put in front of the reception. Correct now? So let us imagine when this reception was being built, ArivuPro was looking at some good paintings. So what did they say? I don't know how many of you know. In Jayanagar, there is something called as auction house. You guys know? In Jayanagar, there is something called as auction house. Weekends, they conduct auction. Anything can be got to the auction. As if, I mean, as long as they are antique items. Telephones will come, the old telephones, like this it was there, no? They will come, gramophones will come, paintings will come. Now, paintings will generally keep coming. So ArivuPro said, sir, can you go and get us the paintings from this place? I said, okay, I will go and get it. What? Paintings. Because I know it is there in the auction. They have put a newspaper advertisement. I'll go and participate in the auction. I said, ArivuPro, I will get these paintings for you, unique paintings for you. Now I have agreed to get it. Tell me what type of goods it is. I have agreed to get these paintings. What type of goods? Ascertained, unascertained, future, contingent, what? What type? Contingent goods. Why? Macha, I can go to auction. I will bid for 2,000. Someone says 10,000. I'll say 12,000. Someone says 1 lakh. I come home. I do not know. Just because I go to an auction house, that doesn't mean that we will pakka get the painting. Auction is a contingent goods. The best example, until IPL, last hammer is dropped. You never know where that player will go. But the players, the owners will go thinking we will get him today. Agreed? No? Yes or no? So remember, auction is always a contingent goods. Agreed? Huh? Hello? Done. Types of delivery. What do you mean by delivery done? Voluntary transfer of possession is called as delivery. Okay. And delivery can be classified into 3 things. One is called as actual delivery, constructive delivery, symbolic delivery. What do you mean by actual? Legs packet, anta, done. Physical delivery of goods to the buyer. Directly I am giving you the goods. If a seller is directly giving the goods to the buyer, it's called as what people actual delivery. The next one is called as what people? Constructive delivery. What do you mean by constructive delivery? So, for example, let us imagine I have parked my car in a second-hand car showroom and I'm selling it. And I've also put a ad on my FB, Facebook and Insta that this car is for sale. Anyone interested can please contact. Someone called me, sir, we want to buy the car. He asked me how much. I said around 7 lakh rupees. He said, sir, can you reduce a little? I'll say, see, 7 is the maximum, but okay, I can go up to 6 lakh rupees. He said, okay, where can I check the car? I say it is here. He said, okay, sir, I'm okay. I'll go ahead. He sent me the advance amount also. Everything is done. I said, okay, sir, you're the owner. Go ahead, done. Now, people, where is the car? The car is not with me, but where is the car? The car is in that garage. Now, what will I tell? I will call that garage person and say, hey, going forward, don't give the car to me. There will be one more person who will come and collect the car. You give the car to him. He'll say, okay, sir. Correct, huh? Did the car move even 1 inch? No. But don't you think delivery was made from me to him? This is called as what? Constructive delivery. In a constructive delivery, there will always be no physical movement of the car or no physical movement of the goods. It will be in someone's possession. They will inform you, acknowledge. That's the word you need to write in the exam. That's the keyword. The garage person acknowledged, okay, sir, I will give it to him. That's all. That is called as delivery. Now, this whole process is called as constructive delivery. When delivery is effected without change in custody, wherever it was, it is there only. But still, delivery is completed. Understood? Hello? Third one, symbolic delivery. What is symbolic delivery? To deliver one thing, we give something else. For example, to deliver a car, what do we deliver? We deliver a key. We call this as what? Symbolic delivery. So if we give the keys, that means we have given the car. Agreed? Yes, sir. That is called as what? Symbolic delivery. Next one, there are two types of documents. One is called as document showing title. Next one is called document of title. What do you mean by document of title? Document of title means, people, the document itself is the ownership. Whoever has this paper, imagine, people, a 100 rupees note has fallen down. It is mine, but whoever picks it, aren't they the owner of it? Correct? The world will tell you, sir, this is not yours, it is that person's. No. Whoever has this document, they itself are the owners. Hello? Best example, bearer instrument, bearer check. Promissory notes, now you would have seen, no, bearer check. Bearer check, name is not there. Whoever finds it are the owners of it. Hello? Correct now? What else can be the example of document of title? Railway certificates, warehouse certificates, war finger certificates, everything is go downs only. For example, imagine you're going for a shopping or a movie. You have to deposit your luggage in front of the theater or in the shopping complex. You have to deliver. You have to give your luggage. If you give your bag, they give you one coupon, token. Now, people, let us imagine you lost that token somewhere. Someone goes and gives that token to the security guard. Will he get the goods or not? He will get. He will not ask for ID card, Aadhaar card and all. Whoever has this token, that person is the owner. Document of title. Hello? Next one is called document showing title. What is my document showing title? Even if you lose the document, nothing will change in your life. Example? Share certificates and any other example. Aadhaar card, your driving license, your bike's RC. Even if you lose it, the person who gets it will not become the owner. Best example can be, imagine you got your CS certificate. You cleared your final. You lose it somewhere. Someone gets it, they'll become CA. Yeah? No. That's what I'm telling you. These are all documents showing title. They are not the owners in its own. Agreed? Hello? Okay. Next one is, people, contract of sale. It can be of two types. One is called sale. Next one is called agreement to sell. Tell me, what do you mean by sale? What is agreement to sell? Sale, ownership is transferred immediately. Agreement to sell will be transferred in the future date after fulfillment of condition. Risk is with whom? In sale. In sale, ownership is transferred immediately. Hence, the risk is also transferred immediately. The risk is with the buyer. Agreement to sell. Kisan company said, we will buy tomatoes after 6 months. Agreement is made today. What if after 3 months some cyclone comes, entire tomato crop is gone? Who will bear the risk? Seller, because the ownership is not yet transferred. Ownership will be transferred only after the contract of sale. Your crop has to come from uncertain goods. It has to become ascertained goods. That's when the ownership will pass. Agreed? Yes, sir. Okay, that is called as sale. That is called as agreement to sell. And there are some differences no in this chapter. What and all? Hire purchase. What is hire purchase? Hire purchase. Hire purchase. Whenever you are buying a product, the possession is transferred on first installment, but the ownership is transferred on the last installment. Such type of contract is called as what? Hire purchase. Correct? What is the in the hire purchase? Risk is with whom? Ownership is with whom? Ownership is with whom? It is with the seller until the last installment is made. So the risk is with whom? Hirer, that is what? Buyer? Seller or hirer? Seller. Ownership is with the seller, correct. But risk is with whom? Buyer or seller? Buyer or seller? Buyer. So buyer or seller? It is with the seller, people. Risk passes with the ownership. Yes or no? Huh?
No such risk.
The owner has?
No such risk.
Which risk?
No risk.
Like I didn't get you.
No such risk.
No. What I'm saying is in hire purchase, who is the owner? Seller. The owner is seller is the owner. So whose risk it is? Anything happens to the product, whose risk? Let us imagine this TV was got on a hire purchase. There's a earthquake that came in between the class. Split, TV went inside, earth came back. Now tell me who will bear the risk? Is it seller or buyer? Seller or buyer? It is seller. In hire purchase, you have a risk. Once again, I'll complete. Seller only is liable. Pakka. But what is the exception? Now, seller's goods are with us. Now, it is my responsibility to take due care of this product. Then, when earthquake is happening, due care means what? I have to hold two earths like this. What due care I will do? So due care means what? It is my duty to check whether have I installed it properly or have I installed it negligently. That risk is on me because it is a contract of bailment. So his product is with me, it is my risk. Understood? Now, sir, what do you mean by? Now I'll come to your point. You said, sir, in hire purchase, owner takes no risk. What do they mean? They mean, what if the buyer becomes insolvent? In such case, what will happen in the case of hire purchase? Because the ownership is not yet passed, he will come, he will uninstall the TV, he will take it and go. That's all. But in sale, what has happened? Ownership is passed. I am the owner of the TV. You cannot come and just let and take it because it is my ownership. In hire purchase, the owner is still with the seller. After repaying the last installment, I will become the owner. Understood? Pakana? Yes, sir. That's why we say in hire purchase, there is no risk. Clear? Okay. And what else is there? Bailment and sale. What is the difference between bailment and sale? Bailment only possession, sale ownership. Bailment can be free even for cash. Sale can never be for free. And in bailment, product is always returned back. In sale, not returned back. Correct? Yes, sir. Sale, hire purchase, agreement to sell. Done. And the last thing in this chapter was what? Ascertainment of a price. Important. How do you ascertain a price? First one, by contract between the parties. Meaning, in the contract itself will say that the price is 10,000, pay 10,000, done. Correct? Next one is a course of dealing between the parties. What do you mean by course of dealing? What is the big difference between these two? Contract is people one time, course of dealing people, repetitive in nature. That time I cannot write the price in the contract. For example, there is a farmer who is supplying, say, fruits and vegetables for some supermarket, Tata supermarket. I'm agreeing for next 2 years I will only supply. But can I write onion will always be 50 kg in contract? Can we write? No, it keeps fluctuating. That's the meaning of course of dealing. That day price we will give. How we will arrive at that day's price we will check. But it cannot be constant. That's the meaning of course of dealing. Clear? Hello. Third one. Whenever there is a contract between seller and buyer, seller has given the possession, but they have not agreed on the price. What to do? No. Seller has given the possession. Buyer has taken the possession, but they have not agreed on the price. Is this contract valid? Is it valid? What's your name? Pramod. Is it valid? Is it valid or not? Price is not agreed, but the product is given. Is the contract valid? Price is not mentioned. They have not discussed at all. Understood? Half of you will write and come. It is uncertain, vague. It is valid, people. Remember, in Sale of Goods Act alone, not in Indian Contract Act, in Sale of Goods Act alone, if at all there is a product, if the product is transferred, I mean the ownership Allah, I'm saying the product, the goods are transferred. The buyer has got the possession and the price is not agreed means you will have to write the buyer has to pay reasonable price to the seller. What is reasonable price is matter of fact. It depends upon the product. But what I need to pay is a reasonable price. Is this clear? Hello? Next one. They can determine the price depending upon a third party that is called as valuers. Now, what do I mean by that? A wants to sell his car to B. Recently, my friend sold the car. Their agreement was simple. They will call the spinny guy. You need to pay, I think, around 1,200 rupees. Spinny guy will do 2 hours of inspection. Literally 2 hours. And you know what? The inspection will never be done in our parking lot. It will be taken to the daylight, meaning they will take it outside. Some 8 to 10 kilometers they will drive. They will park wherever there is sun. They will not do inspection post 6 o'clock. And even I was shocked looking at all of that. And he has easily clicked around 180 to 190 pictures. He will go underneath the car, he will click there, he'll open the bonnet, click there, every 180 to 190 pictures he has clicked. So, so what did these two people agree? A and B. Macha, we will sell the car. I am saying 10 lakh. You are asking for 1 lakh. Why risk? If you still want to buy the car, we will call the spinny guy. Whatever he says, we will sell it at that price. He will evaluate everything. He will say the price of this car can be somewhere between 5.5 lakh to 6.25 lakh. Now the buyer will ask for this price, seller will ask for this price. They will settle at this price. Correct? Yes, sir. Now this is only called as what? Third party. Agreed? Sir, let us. Now what happened? A and B, today they saw the inspection. They will take around 1 day to give you a detailed report. So A saw the car and he liked it. A said, okay, let him give a quotation. I will start using the car. A has taken the car also. Yes, sir. Okay, sir. Sorry, B has taken the car. He started using it. Before the report came, he started using it also. Now, people, the spinny guy was not able to give the report. Something went wrong. He was not able to ascertain the price. Now, in that case, what to do? Should I avoid the contract?
Avoid, sir. What because you have agreed with, sorry, he has not given
The buyer should
the
receive the
contract.
So, if at all the buyer has not received the goods, you guys will avoid the contract. If the goods are transferred, if the goods are already received by the buyer, then what you will pay is reasonable price. Remember, exam point of view, very important. Pakka, there will be a question. Again, I repeat, whenever you are agreeing that third party will evaluate and give the price, and if third party has evaluated, but he was not able to give the price because of any reason, but the goods were transferred to the buyer. Now the buyer's responsibility is to pay whatever is a reasonable price to the seller. Then the goods are not transferred. Yes, the contract can be avoided. Void. Clear? Hello? Yes, done. Next unit, sir, unit 2, conditions and warranties. Now, what do you mean by conditions and warranties? Whenever there is a sale from a seller to a buyer, the seller will make hundreds of promises to sell his product. All these promises can be called as statements. These statements in this chapter can be called as stipulations. The promises made by the seller to the buyer at the time of contract of sale is called as stipulations. Some promises are very important. Some promises are okay. You can ignore them. The promises are which are very important. Upon that only the contract is standing. We call that as what people? Conditions. The contract is depending upon the very main thing that is called as condition. If that is not met, the contract only is based. Whereas the other part, you have made some promises, but they are not very essential. Then you will call it as what? Warranties. For example, sir, Nitish will go to a shop and say, I'm going to Kashmir. I want a jacket which can withstand the weather conditions of Kashmir. Now the sales guy will give him a jacket. Now Nitish will believe in him. And he'll say, is this good enough? He says, yes, it is good enough. Now they take it. Now he goes to Kashmir. But when he is wearing that, people, it is nowhere taking that cold of Kashmir. He's not able to withstand that temperature. Now the question is, there is a promise made to the shopkeeper, sir, this is a very good product. It can withstand Kashmir and you go to moon only. Why astronaut suit and all? In fact, NASA approached us for this suit. Yeah, now they will promote so much. They will promise everything. Now, don't you think the entire contract is standing on a main element that it has to withstand the cold weather? Now, if that does not satisfy people, the contract can be avoided. Nitish can use it there for 7 days. Not use it. Simply is that it is your duty to come and give back the product. You can claim back your money along with compensation. So, cabinet tempter very good. Now, how do you expect him to try it? Sit in fridge. That's what I'm saying. How do you test? So, if it is okay, I'll give you to like this. If you no, 1 second. Have you purchased any raincoats? Have you tried it? Why? Then why do you expect him to go and sit in fridge? See, you believe that the product works. You go to a product. I believe all of you would have done. They sell it as raincoat. You buy it. Now, if it is not stopping rain means, agreed, no? Other, that is what the main essential element is there. What raincoat? Why do we wear? It looks cool. Hoodie and all comes. No. So KVA tempter 100% true. What is it is true, but it depends upon. In KVA tempter only, there is something called as quality or fitness. When the buyer has made his purpose known to the seller and relied upon the decision of the seller, then the seller is liable. Quality or fitness, implied condition. Hello? Understood? Fakana? Okay, so whatever conditions are important, they are called as, whatever statements that are important, they are called as conditions. Remember, if conditions are not met, breach of condition, then what will happen? Breach of condition will give you a right to cancel the contract, give back the goods, get back the money. Plus, you can also claim compensation. Sir, warranty. Warranty is what? He got the jacket, but probably some 2 stitches are open here, or something like that. Probably one button is missing, which is ignorable. If that is the case, then yes, people, he can get it repaired. Go back, ask them to fix it, but don't even give extra 1 rupee. That is called as what? Warranties, which is not essential to the contract. Hello? Pakam? Okay. Next one, sir. When can the breach of condition be treated as breach of warranty? When can we do it? First one, when buyer waives off stipulation. What do you mean by buyer waives off stipulation? Nothing but people, we all fall here only, give up. You guys would have purchased the product. You know that it does not fit your purpose. What do? You give up and you come. Correct? Huh? In that case, you have a right to go and give back the product. What did you do? You did not give it. You adjust it. That is only called as what people give a waiver. Next one, treats breach of condition as breach of warranty. What do you mean by that? A ordered 10 kgs of basmati rice. Yes, sir. Meaning, let us imagine basmati beda. I have ordered first grade of quality rice, first grade quality, which is around 100 rupees per kg. Now, people, what was delivered to me was second grade quality of rice, which comes around 70 rupees per kg. Don't you think in these two contracts, the main essential element is the grade, the quality of rice? The entire contract is revolving around quality of rice. So I ordered this, but I got this. Now Nitish ordered this. Nitish cooked biryani. Nitish fell in love with this rice. Wow. Now Nitish said, why not grade 1? Grade 2 only is good. He is convinced. Now what is he doing? He has a rights. I mean, he has right to go and give back the goods because the main condition was grade 1. That's why I paid extra. Hello. I have a right to go and give it back. But what did Nitish chose to do? I will not give it a macha. I will accept it, but not like condition 1. First one I gave up. In second one, I will not give up. I will at least go and get back the extra money I have paid. 30 rupees I will go and get back. Hello. Second one. Understood? Treats breach of condition as breach of warranty. Contract is non-severable and buyer accepted it. What do you mean by this? Contract is non-severable, buyer accepted it. Nitish got his jacket. It did not serve its purpose. Breach of condition, but Nitish liked the look and feel of it. And it is reversible. You wear like this, you wear like this. Every way it is working. Nitish is impressed. Now, people, I cannot separate it. It is not serving a purpose also, but I like the touch and feel and look of it also. So, Nitish compromises and decides to keep it. And that is what is the third condition. What? Contract is non-severable and buyer accepts it as a whole. Hello? Okay, the fourth condition, fulfillment is excused by law. This is nothing but what people? Supervening impossibility or why did you not, why were you not able to complete the contract? The reason is because of change of law, change of circumstance. Because of that, I was not able to complete the contract. So that means what? You cannot claim compensation. Why did the other party? In our question also we saw, no. What is that? What is the compensation he can claim? We saw that question, no. No, not that one. The water something we saw. 750 rupees. So why did I not do it? The Apple thing, right? Was that question we saw? Not that 700 rupees, 750 rupees, and 500 rupees. Ordinary and special. Why was he not able to deliver? Correct? The contract, why did I not perform? Because not of my fault. There is something not in my hand. That is the meaning of excuse by law. Imagine COVID, lockdown, alien enemy. Now, in these cases, I cannot perform. You cannot claim compensation. Whatever you have given me, I will give back the money, but I will not be liable to pay compensation because it is excused by law. Law only is telling me, give back the money and be done with it. Do you need not have to pay compensation and all? Law only said, then okay, I don't have a problem. Understood the four scenarios? When the breach of contract will be treated as breach of condition will be treated as breach of warranty. Clear? Okay, next one. There are two types of stipulation. One is called express, whatever you guys have agreed. Next one is called implied. This is something which you have not agreed, but law says it is still to be there. The stipulation implied can be further classified into implied condition, implied warranty. That means what? This is something which you guys have not agreed, but it is still there in the contract. Hello? Okay. Now, implied condition. The first one is called as implied condition as to the title. For example, people, yesterday I said, I'm selling you the mobile. Correct? Now, whenever such things can happen, whenever you're buying something from any shop, or on street side, anyone shops, anyone purchases? No one? All yellow. No. Street side we purchase. We get all nice clothes and all, shoes and all we get it. Yes or no? Da? Now, are you sure that shoes is brand new? Boys, I think you can relate to branded shoes and all you will get. I tell you where you will get also. There is one very famous bazaar on it. Chor Sida, how popular it should be. Alas, look at the country. India is not for beginners. Chor Bazaar, everyone knows that it is not fake. Legally, they are doing illegal system. Change the name only. And sad part is, it is there in the map as Chor Bazaar. Chor Bazaar is, it's not something it is known. It's a landmark. So wherever you go, they put there. Even if it's selected, it's there in multiple places. Delhi, it's there. Pondi, it's there. Yeah. Now tell me, you go there, you buy it. You ask them, Anna, this is yours only, yeah? But technically, you tell me, is it theirs? Implied condition. When a seller is selling the goods, you will not ask, Anna, is this yours? You will not ask. But it is an implied condition that it will belong to him only. It's assumed. But what if that is not the case? What will you do? Imagine we purchase something. Now someone comes and says, Nitish purchased not shoe. Jiva comes and says, hey, that is mine, special edition. No, see, I have signed it here. On the sole, he has signed it. Now tell me, what should Nitish do? Nitish can use it. Nitish has to give it back. He can give that shoe alone.
He can get the compensation from sales.
But compensation is okay. Tell me what to do with the shoes. Can he keep it or should he give it back? Original owner, he has to give it back. Remember, people, giving back the goods is mandatory. Nemo that quod non habet. No one can give what he does not have. If I am not the owner, I cannot give you the ownership. So it is your duty to give it back to the rightful owner. Hello. Yes, you can claim compensation and all, but what to do with the goods? You have to give it back. Question can be asked on that part. Remember. Next one, description. What do you mean by sale of goods by description? Nothing but something which describes the characteristic of goods. Basmati rice, fresh sweets, anything which is describing that particular product. That product has to meet that description. Mysore silk, Kanchipuram silk. I don't know what else, something else. Mysore peda, Mysore pak. Correct, whatever. So these things are called as what? These things are called as description. You have to meet Tirupati Laduna. Okay, maybe. Yeah. So that is, you have to meet that description. If description is not met, correct, everything. Assam tea, Darjeeling tea, Ooty and all. Correct. Uh-huh. They sell, no. No, they sell it in few places. Huh? No. Let us imagine you give me money and say I'll get you Tirupati Laddu. What if I give you some other Laddu? Huh? Correct? No. Now, people, let us imagine. If at all your now imagine they sell something as Assam tea. Hey, how will you know the Assam tea? Then Assam tea will be orange in color. That will also be same in color. How will you know? Exactly. On packet only they're telling you Assam tea. What is the guarantee? Huh? Exactly my point. What is the guarantee? To print, I will print. FSSCI. Maggie ate. Huh? For 2 generations we ate. FSSCI.
GST. That number, sir.
Holy bro.
Sir, active will happen, sir.
Okay. It's that. Holy bro. Understood now? So in simple, as a seller, I need to make sure it is an Assam tea. It has to be a Darjeeling tea. Buyer does not know how to get it, but you cannot cheat it and you cannot take more money by adding that word, because by adding that word it gets sold. I cannot take advantage of it. That's the meaning of it. Next one, sample. Sample means what? Again, you go to a shop, they will give you, especially I tell you, dry fruits. If you go to a mall, they would have put everything in jar. I taste there, different. I get it at home, different. I don't know why. There it will be very nice. In home it will be waste. It happens, in many cases it happens like that. Especially I'll tell you, nowadays it happens or not, I don't know. Now they will have some, this market where they'll be showing some like equipment, gadgets, tools, like vegetable chopper. They will do, hey, sir, see, you can use it at no, I go and do, not even once it will work. Huh? That Mosambি thing used to come like a pipe. If you put it, juice will come. Yeah, juice, nothing can. 2 times, third time it will break. That is what is sample. All kaldro, chor. They will show this. But the bulk will not correspond to that. That is exactly this point. That is, if you show something, whatever I'm selling, both has to be same. That is what is the meaning of sample, correct? Next one, sale by sample and description. What do you mean by sale by sample and description? Have to meet with the sample also, have to meet with description also. So I show basmati rice in a cup, and that basmati rice, whatever is shown in the cup, that should also be matched. And also a tag called basmati, that should also match. Next one is quality or fitness. Nitish goes to the shop. He says, I want to buy the jacket fit for Kashmir. I have made known my purpose. I believe in the seller's choice. I believe in the seller's decision. And if that purpose is not served, I have a right to give back the product, get back the money. But remember, people, if at all the product has single use, you need not even tell the purpose. I will take it home. But if the purpose is not served, I can come and give back the product, take back the money. Example, this is where you guys saw the case of, what is that? Kettle hot water.
Yes, sir.
Mauli? Yeah, Guru. Handy versus backside. Priest versus last. So in this case, what happened? They poured hot water into one. So a person went and purchased the what do you call that, flask. He purchased the flask. He went home. He poured hot water into it. He closed the lid. He gave it to his wife. The hot water, that is flask, became an atom bomb. Blasted. The person, what did he do immediately? He did not go to hospital. He went to the shop first. Money important. He said, hey, bomb blast happened. Now people tell me, is he liable? Let us imagine. He did not say, give me the flask and all. Remember, flask has a single purpose. It is made to put hot water. Because if not, why will I buy that? I will buy normal bottle. Don't tell me, sir, you can put normal water also into it. Then that is the case, I'll buy normal bottle. I'll not, why will I pay extra money? Hello? Agreed? So single purpose, even if I do not communicate, I will be liable. Example for any product having multiple purpose. Rope. Rope can be used for what? To hang clothes, to hang. Mean multiple purpose. Correct? No. So now imagine you asked rope, he gave it. He thought you are using it for hanging the clothes. You are using to swing hang alla. Very adharale. Now people, now I have made known the purpose. The product has multiple uses. In such case, people, I will not be liable. Hello? Done. Remember people, this condition will not apply in the case of products purchased under trademark. Why? You go to a shop. Imagine you go to some big mart. There are so many branded shoes. The salesman will not say anything. You will go and pick up the brand you guys want. It can be Adidas. Very less amount of effort is put by a salesperson. You made your call because the brand called you, not the sales guy. That's why if at all a product is purchased under a trademark or a patent name, this condition will not apply. Hello? Okay. Merchantability means what? The product has to be free from defects. But remember, this is subjected to caveat emptor. You go and you pick up something which has defects, it is your problem. Agreed? Last one is called as people wholesome. What do you mean by wholesome? Wholesome applies in the case of edible items, perishable items. If I purchase sweets, it should be fresh, bread, fresh. It should not be stale. That's the meaning of it. Clear? Hello? Okay. Okay, let us do one thing. Let us end up here. At 4:15, they have a different class. I think students have already sat there. I know. Even I'm irritated what to do. Because it will take time for them to set up and all of that. Let us catch up tomorrow. We have to. Okay, we'll do it. Huh? I could have completed this part, no? It will take 15 minutes at least. Let me not just rush it up. It's okay. Done. Chalo, thank you all. See you tomorrow. Bye-bye. And tomorrow we'll do more questions. With whatever units we have done, read and come, we'll do questions tomorrow. See you. Bye-bye.
Okay. So we were doing implied conditions and implied warranty. We had done implied condition as per the title. What do you mean by that? A person who is selling the product, we believe that he has the ownership, or a person who has agreed to sell the product. We believe that on the date of sale, he will have the ownership. Description is whenever you are selling a product with any characteristic attached, Assam tea, fresh sweets, these are the questions that will come also. Yeah. So for example, one question had come. A seller sold certain sweets saying that they are fresh. And he gave that sweet as a sample also to the customer to taste. When tasted, it was really good. So he purchased 1 kg of sweets. He went home. When he saw the sweets at home, the sweets were spoiled. So they're asking you, does the customer has any redressal remedy in this particular case? Does he have? What is the remedy? What is the provision? Sale by sample and description. Because it is met with sample. That is, I mean, it comes with both. You're saying it's fresh sweets. It has to be fresh. And sample I tasted did not correspond to the bulk. Yes. So again and again and again, I'm telling you, start using these words in the exam. Hello. Okay. Next, sale by sample and description. That is what it was. Quality or fitness, we saw Nitish case. Quality or fitness, what did we see?
We should definitely test the purpose and say.
The buyer has to convey the purpose.
Yes, all is
He relies upon the seller's skill and judgment, and buyer must have relied upon the seller's skill and judgment, and seller should be of the same business in the ordinary course of business. Okay, in such cases, then whatever KVA tempter also will not apply. Your jacket case, KVA tempter will not apply. Okay, in this case, now what is that they're telling you? Whenever there is single use, then if the product has only single use, I did not communicate my purpose. When the product has single use, there is no need to communicate the purpose. Example we saw was the same flask, correct? Next was if there is a patent or a product purchased under a trademark, what will happen? Seller is not liable. Agreed? That is where, and we saw merchantability and wholesome. What do you mean merchantability? Free from defects. Wholesome means it has to be, in the case of perishable and edible items, it has to be free from defects. It should be fresh. Okay. Yes, yes. Anything which is perishable and edible, fruits, vegetables, milk, these are the examples they ask you as well. And one more thing also, the sweets example. Why does it come under wholesome? I just now gave the example, no? Why should I write it in a sale and description? Why not wholesome edible, right? Again, I tell you, hint in exam for a reason they told you. He claimed it as fresh sweets. He gave it to you to taste. This and all simply they'll not tell. There will be a reason. That's why I tell you always, you will be smart if you know the hint. Every question will have a hint, and you know that hint is nothing but it will be there in your provision. Those words will be there in the provision. That's how you need to pick it up. Yes. Yesterday, someone was asking, what is the activity we can do to improve our provision of law? See a question, take a book, read the question, don't write the whole answer. Just write the provision of law. Now, I told you one question. Don't tell me from head to toe. See, for writing practice, have 3 questions a day. For provision practice, go through the question. In one place, keep writing the provision. Now, I told you this one. Sale by sample and description. Done. That means you know how to present this answer. If you are not getting that, you don't know. Go and read that. The more you do, the better for you. Hello.
Yes, sir.
Okay. Next one, people. Implied warranty. Share YouTube link. Which one? Bangal Mangari. Which YouTube link I should share? Okay. Implied warranty. Warranty has to undisturbed possession. Yesterday, we sold Nitish's phone. I gave it off to you. You tell me from tomorrow what will be your life. Nitish will come every day, early morning. Hey, give me my phone. It is my phone. Evening again he'll come. Night again he'll come. Technically, I have sold it to you. You are the owner. But every day someone is coming and disturbing you. They please give back my phone. As an owner, is that the way you want to enjoy your product? Answer is no. That's the meaning of what? You have a right to enjoy the quiet possession of the product. Undisturbed means what? There should be not anyone coming and asking for the product, claiming that it is mine. That's my right to enjoy a quiet possession. If I have to tell you the other way, let us imagine this way. I've taken a phone, but on a EMI. Now I sell my phone on OLX. I have sold it. Papa, that fellow doesn't know. The bank people have started asking him now. If you don't pay, I will come and take back the phone. Now he is worried. I paid. He has paid complete money and he has purchased the phone from me on OLX. But I've taken that phone on EMI basis. Now you tell me, whoever purchased it, every day someone will keep coming and disturbing him. If you don't pay, I will take off the phone. If you don't pay, I will take off the phone. With that fear, now how will I enjoy the possession of the product I purchased? So that is what is these two things. Non-existence of encumbrance. Encumbrance means what? There should not be any charge, pledge, mortgages, hypothecations on the product, which is unaware. Or disclose it and sell. That's a different story. Do not keep it silent. It is your duty to disclose as a seller. Sir, this phone is on EMI. I've paid 3 EMIs. You need to pay another 6 EMIs. Please keep it in your mind. I have to disclose and sell. I cannot keep it silent. Clear? If I don't disclose, what will happen? Someone will keep going and bothering him. That time, this will breach. Warranty has to undisturbed possession. Sir, now if a bank fellow goes and keeps asking him for money, what should he do? He has two options. One, he can only pay the entire money to the bank, recover it from that seller. Option two, push the seller to pay the money to the ICICI bank, meaning the first buyer, the first person is there, no owner. Tell him, I have paid the entire money to you. It is your duty to pay to the bank. Push him, or you pay and recover it. Exam, they can ask you a question. What are the remedies he has? Remember and go. The little turn on AC, it's completely off. Check if Priyanka is here. She's up. Priyanka, can you check? Turn on AC. It's off. It's on. No, they would have turned off. Last bench fellows. Simply that. See, it is tradition that to blame the last bench. I can't break the tradition and all. When we were there, they blamed us. It's on. Temperature? See, everyone has, that's manipulated. Wait. 25 yeah. 24 ಮಾಡಕ್ಕಾಗತ್ತಾ ಅಥವಾ ಅದು ಫ್ಯಾನ್ ಮೋಡಲ್ ಇದೆಯಾ AC ಮೋಡಲ್ ಇದೆಯಾ ನೋಡಿ ಫ್ಯಾನ್ ಮೋಡಲ್ ಇದೆಯಾ ಫ್ಯಾನ್ ಮೋಡಲ್ ಇತ್ತಾ ಅಲ್ವಾ ದಟ್ಟಾಟ 6 ಟೈಪ್ ಟ್ಯೂಬ್ಲೈಟ್ ಮೇಲೆ ಇಟ್ಬಿಟ್ಟು ದಟ್ಟಾಟ ಅಂದ್ರೆ ಓವೆನ್ look at the light that comes. Okay, see here. Non-existence of encumbrance is clear. Hello? Quality or fitness by usage of trader. What do you mean quality or fitness by usage of trader? For a particular product with over a period of time, it would have been accepted to use that product in a particular way. For example, if I give you a pen, what will you use the pen for? Depends, sir. If munde around irritate, will keep like this, sir. So, you know that the pen is used for a particular purpose. But if you are deviating as a seller, I have designed a pen, but which is not fit for writing. It is my duty to disclose that, sir, traditionally this product was serving this purpose. Today it does not serve that purpose. It is my duty to disclose. Now, for example, one example I can give you is, I would have given you that example in your class. Now, if you look at this particular brand, now what is this particular brand? There are two products, two brands. One is called Gucci, one is called Adidas. What did they do? They have come up with the umbrella. Yesterday he said no, raincoat. Correct, no? Now see, they have done one umbrella. What do? You purchase that umbrella. What is the umbrella used for? Rain, no. Now you will also believe it by no, you will test. There only, Anna, ಸ್ವಲ್ಪ ನೀರ್ ಹಾಕಿ You will not test, no. Agreed or not? And that to imagine, what is the price we pay for umbrella? 1,000, 500? Yes, to something, one amount is there. Will not pay beyond that. Now, what will be your feeling if you have paid 1 lakh? So you expect it to stop even thunderstorm also. Lighting it also, it should stop. That is what will be your expectation. Now, people imagine Gucci and Adidas has come with the product. 1 lakh rupees is the umbrella. Traditionally, umbrella is used to stop rain. But this will not stop rain. Eppadi twist? This will not stop rain. See, they will keep in temple for God. This is the answer I was looking for. What did they design it? To keep it in temple for God. Correct. So, people, why did they design this? They designed this people as a part of interior decor, sun protection Allah. They have given, if you go and check their website, they say the purpose of this is as an interior decor. Hey, who will take this for Sunday? I mean, so of course, they say that it does not stop rain. We take it outside. So if you check their website, they say that it's a matter of status as an interior decor. Ali was moole see fact there. Open and keep it in one moole. Vastu. Yes, sir. Now, traditionally, umbrella is used for what purpose? They are telling you then when you're selling it in your shop, up put one board. It's an umbrella, but which will not serve the purpose of stopping rain. This is the meaning of quality or fitness. Fitness here means what? That product has been used for stopping rain over a period of time. Now you are deviating it. Very good, creative guy. But you have to disclose it and sell. You cannot keep it silent. That is what is called implied warranty. What is the difference between implied condition and implied warranty? Implied condition also quality fitness came. Here also quality fitness came. There, the buyer has made the purpose known. I have told why I want it. Here, I have not said nothing. Traditionally, you guys shop a lot of things. Why? Because it has been used for a particular purpose over a period of time. It has to serve that purpose. Hello? Pakka? Okay. Next one, people, is called disclosure of dangerous nature of goods. What is dangerous nature of goods? If at all I'm selling you something, people, if at all there are any side effects because of that, it is my duty to disclose when I'm selling it. Best example is if I'm selling you perfume, I have to disclose that it is highly inflammable. If I'm selling you cancer, Mukesh, ad comes no. Yes or no? And whatever is the nature, we have seen it, right? Whatever you are selling the goods, if it has any dangerous nature involved, it is a duty of the seller to disclose. If you don't disclose and sell people, I will be entitled for the damages. That's what they're telling you. Clear up? Hello. Last one, sir, is KVA tempter. Now, what do you mean by KVA tempter? Let the buyer be aware. That means what? The law is trying to protect the seller always under KVA tempter. Agreed? When I say let the buyer be aware, that means what? I'm protecting the seller. You know the opposite of KVA tempter? KVA? Send it or KVA vendor. It's called vendor. It's not there for us, just telling it for your information. Let the seller be aware is called as KVA vendor. Now, what are they trying to tell you? Let the buyer be aware. Exceptions to let the buyer be aware means we are trying to still protect the buyer only. KVA tempter, we are protecting seller. Exceptions to KVA tempter, we are protecting the buyer. What is the scenario? Whatever we have seen in the top. First one, fitness or quality or usage. What is this? When I have made my purpose known. Last case, I have relied upon your judgment. Now, I will not check your jacket. I'm not expecting you to go and sit in the fridge. Don't check. It's okay. It has to serve the purpose. Hello? Goods purchased under patent or brand name. I would have told you in the class. What did we see in implied condition? Whenever goods are purchased under patent or brand name, is seller responsible or buyer responsible? Buyer is responsible. Then why is it coming under exception here? No, remember, under the explanation, they have still given the same thing. It's a wrong heading here, that's all. You have to write it under the exception, but still, who will be protector? They will protect the seller only here, not the buyer. That's how the explanation is also written. If you ask me, it's a wrong classification. It will not come here. Clear, huh? Third one, goods sold by description. Upper we saw Assam tea. I cannot go and check in Assam and see, oh, this is how the leaves are. I will not know. You tell it as Assam tea. I believe it as Assam tea. Next one is merchantable quality. Amazon ta bacha. When you're getting phone on Amazon, you take me only. How unlucky I'll be. I purchased one phone. Yes, sir. Even I did not check. There is this, you don't know, no, that Flipkart, Amazon, and all. You have to give that OTP when your unbox is doing. I checked everything. I gave OTP. After event, I went for that scratch guard where that screen guard you have to put. That time he's telling, sir, see in the center there is one scratcher. Screen center there will be one scratcher, which is not evident at all. OTP is given. Then what else I can do? Done. I could not return. Same mobile I'm using. Where did I return? That's all. If you miss on that day, you cannot return it. I'm saying I just checked it within one day. Merchantable quality means what? It will be free from defects. Sir, now yours had defects. No, that's why whenever the goods are sold by sample or merchantable quality, you should be given an opportunity to inspect the goods. It was given. I did not inspect properly. Done. I can't do anything. Literally can't do anything. Understood? Yes, sir. So merchantable quality means it has to be free from defects. Caveat emptor, I have to check it. But law will protect me. Amazon, law will still protect me because I was not there at the time of sale. OTP, every place they tried to protect me. But still you don't know how lucky we are. Yes or no? I am full lucky fellow. My luck will be, you don't even ask. Literally, I'm lucky. So in Sri Lanka, there is one place. Everyone will go in a train thing. It's very popular, it seems. So we also booked everything is done. It's called Candy to Ella. That's the place. The train journey is beautiful. Like it goes under tea estates, full nature, 7 hours of drive. Beautiful. I did not get the ticket. I tried black, influencer, nothing I got. Okay. Why? Because the entire world goes from Candy to Ella. Now what did I do? I tried the other way. Ella to Candy. Route is same. It's okay. So my entire itinerary. So see, the world will go to check. I mean, to go. They go to Sri Lanka in this way. Now because this one ticket I did not get. What did I do? I had to go this way. So I did so much of Tyaga. So much of Tyaga. So I reached Ella also on time. Tomorrow is my train. I'm telling you 1 week back instead. Tomorrow is my train. Today, people, that entire route, landslide. Full track only is damaged. Guttala, that is how lucky I am. This is how my luck will be. ಹೆಂಗ್ ಬಂದ್ರ ನಾನ್ ಟ್ರೈನ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಕ್ಯಾಬ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದೆ ಇನ್ನೇನ್ ಹೆಂಗ್ ಬಂದೆ I came in cab. I was not in train. So what I said myself, I'm so lucky that luckily I was not in train at least. They like this, there are so many things done. This is one now. For example, I think I would have told you also. I went once to Taj Mahal. You know, beautiful and all. When I went to Taj Mahal there was renovation. The sticks. You imagine seeing a building with sticks, how it will be. I'm saying at least 100 sticks were there when I went. 100 sticks. I just told myself, I opened Google, same. I came back. That's all lucky I am. Every place like this only. Nice, no? Okay. Sale by sample. Sale and description. Sample by description. Sample and description, whatever we saw. The sweets. So if it does not meet to the description or to the sample, you are liable. Trade usage, umbrella. Seller actively conceals a defect, nothing but fraud. The contract is avoidable and I can also claim damages from you. Then, okay, third one, transfer of ownership and delivery of goods. Always remember the primary rule, the risk always transfers where? Ownership. Now, it depends upon what type of goods it is. Because we know there are so many types of goods, existing goods, future goods, contingent goods, uncertain goods. In all these cases, when is the ownership transferring? Because it is very important to know. Now, for understanding that, they're telling you it depends upon the types of goods. Depending upon the types of goods, it can also be decided when the ownership will pass. If it is goods in deliverable state, what do you mean by goods in deliverable state? Everything is ready. Everything, literally everything is ready. Now, when will the ownership pass? The ownership will pass when the contract is made. When the goods are in deliverable state, the ownership will pass when the contract is made. Now, what do you mean by that? Now, for example, I go to a shop. I ask for a lace packet, which is there right in front of me. I tear it. I keep it on the counter. I say, I want this. He will take 5 rupees. Now, when the goods are existing, the goods are in deliverable state, meaning I don't have to do anything to this lace. The ownership will pass the moment the contract is made. What do you mean by the contract is made? Offer plus acceptance. Remember, delivery and the payment is irrespective. What do I mean by that? For example, a case that can be built. I'm telling you people, this is little hard to digest because this is what is written in law. But in real life, we follow different thing. Again, I tell you, Indian Contract Act, Sale of Goods Act will apply only when the private agreement is silent. When your private agreements are clear, this particular act will not apply. For example, there is a building called Nexa here. I mean, the corner. Yeah. So probably last year, what happened? There was a rooftop. There was one. What is it? Or a cafe sort of thing. So there was a blast, cylinder blast that took place in that cafe on the rooftop. So the debris, whatever, the cylinder, the roof, it started flying from the top. You can imagine there is I'm not building up, it is real. You can go and check it. There was a cylinder blast. So of course there is a car showroom in the basement. There are cars lined up for delivery. Imagine there are people who are supposed to come and take it, handshake, key, pose. Now, on one of the car, there are some debris of proof which came and fell. That car is already registered in one person's name. He has to come and collect it. Now, the question is, who will bear the risk? In all the records, that car is already registered in your name. Again, sir, take and give another car. The chassis, so engine number will all be registered in your name, and RC will be generated with this particular thing. You have not purchased something, one toy car in everything will be in your name. It's not like, okay, sir, take this car today. That's all. Now you tell me who will bear the risk? Buyer or seller? Macha, in real also, it is buyer only. Maximum what we will do? Seller, because of what else you will do? Now what will the seller do? Sir, engine will be same. I will just check. Did anything happen to engine? No. Then what will I do? I will replace the body and give. But it's the same car. Lifelong you should be thinking like me only. I saw Taj Mahal with sticks. On this car only the debris fell. You have to keep telling it for you. You don't have a choice. What else you do? Because ownership is transferred. The goods are in deliverable state. Hello? What else you will do? The seller can maximum compensate you. Contract will not be cancelled. Cannot be cancelled. Hello? Agreed, huh? Goods in deliverable state. Ownership passes when contract is made. Now you tell me. Delivery is made, huh? Illa. Money is fully paid, huh? Illa. EMIs, then where is ownership dependent upon your money or delivery? Correct only, no?
Other products, it is difficult to digest. This is you can understand. And then, understand, understood, Next one, the goods which are to be put in deliverable state. What do you mean by that? I go to a cake shop. Anna, எனக்கு இது flavor தான் chahiye. I take that cake. He say, Ida madam. So I say, yes sir, idida. Now people, you have selected the cake you want while he was showing it to you. Apdida, it fell landslide. So it fell people. Now the question is, who will bear the risk? Seller, goods are identified. I asked how much is this cake cost? He said, say 1,000 rupees. I said, okay. Sir, idda flavor. When did you make it? 5 days back. Then idda chahiye. Correct, no? Yes or no? We picked that only. Now, he showed it. Contract is made. I asked, sir, can you sell this to me? He said, yes, yes, I'll give you this only, which has been in display for last 5 days. Now, he showed it fell. Who will bear the risk? Seller or buyer? Seller or buyer? So remember people, in cakes, there is one thing that is to be done. What? The goods are in deliverable state. But can I take the cake like that only? No. He will take it. He will keep it. He will write something there. One paragraph. Happy birthday, macha. They should write no. Is it written? The goods are not yet put into deliverable state. Product is ready, but you will not pick the cake like that only. There is something yet to be done. Ownership will transfer only after that thing is done. What is that? Happy birthday, macha. That has to be written. Hello? So what do you mean by goods are to be put in deliverable state? At certain times, the products will be ready, but the fine touch, the last moment thing is yet to be done. Sir, another example, you go into a shopping complex. There is that belt stand where hundreds of belt will be put. What do? You pick the one you want. Agreed? Now you try to put it on. Definitely not our size. Now we will go and say, Anna, please, can you make it to my size? He will take one buckle thing. He will press that buckle. Now we have identified what is there in the belt to be done. It is already in deliverable state. But people, it is not fitting your size. There is something to be done. That is what is called the goods to be put in deliverable state. It is existing, but last second thing is to be done. Ownership will pass only after that is done. Hello? Now, for example, it can be your, say, pant. Your pant is really, you go to, a branded shop. The last part of the pants, they will alter it for you right in the showroom. It can be fit, it can be made fit to your size. Now you pick the pant, in delivery, I mean, the goods are ready. I identify, billing, everything is done. But he will say, sir, do one thing, come back tomorrow. I will stitch it and keep it for you. Now I said, okay. Now I've paid the money also. 9 people, the entire showroom, there is a short circuit. Entire pant is gone, including yours. Now you tell me, who will bear the risk for this pant? Seller or buyer? Seller or buyer? I've paid money also. In car case, you said buyer. That time also seller only. It's not delivered. No. That's what I'm saying. Transfer of ownership has nothing to do with money and delivery. So whether the product is delivered or not, it has nowhere relation with the ownership. Now in this case, what they're telling you, the product is identified, correct? The product is also, you said that you have to put it into deliverable state. What do you mean by that? The ownership will pass only when the stitching is done. The product is now complete. Now there is still one more thing pending. What is that? You have to inform to the buyer. Sir, your product is now ready. Come and pick it up. If it is not informed, the ownership does not pass. Ownership will pass only after that call or information that your product is ready. Hello? Understood? Okay, next one. Goods in deliverable state.
seller has to do something to ascertain the price. Now, what do you mean by this, people? Nothing but the goods are ready. For example, you go to a shopping mart, there are these rice or dal, whatever you guys want to do it, it's there, existing. You put whatever you want, you put it in a packet. The goods are identified. It was unascertained. You have made it ascertained now. When will the ownership pass? They're telling you the seller has to do something to ascertain the price. Now, what do you mean by ascertain the price? Ascertain the price means people have to do something to check. It can be weighing, measure, number. So I have to do something here. Only after that the ownership will pass. That's what they're telling you. Seller has to do something to ascertain the price means the product is identified, but I don't know the quantity. I don't know the number. I don't know the measurement. Imagine you go to you go to buy a you know stitching fabric. You go and buy whatever. It can be shirt, kurtas, whatever you buy. You buy that fabric. Now you go and select the fabric. Now you identify the fabric you want. The goods are identified, ascertained, but you do not know the length you want. The ownership will pass only after seller has to do something to ascertain the price that can be measured. He can say 1 meter, 2 meter, whatever they say. Only after doing that is when the ownership will pass. The question can come. You go to a shop, you identify a garment. Imagine it, you can identify one textile, a shirt piece. You keep it. It is kept on the table. So the goods are identified. Someone spills a coffee over it. Who will bear the risk? Is it on the seller or the buyer? You will write it under this thing. The goods are identified. It is existing. But the seller has to do something to ascertain the price. What the entire bundle I cannot pay. How much would I pay? Correct, right? So that is what I'm saying. After the price is ascertained is when the ownership is passed, is what they're telling you. Understood? Hello. Last one, sir. I mean, sorry, unascertained or future goods. When will the ownership pass? When the goods are ascertained. So when the goods are in bulk, first it has to be separated. Who should separate it?
Is the consent of seller or seller with the consent of buyer?
So who will separate it, people? It will be either the buyer who will separate it or the seller who will separate it. If the buyer is separating it, it should be with the consent of the seller. If the seller who is separating the goods, it should be with the consent of buyer. For example, what do I mean by that? If I go and try to choose some, say for example, I go to buy some tomatoes on street. There is a person who is selling, there's a heap of tomatoes. Now, there are two ways it is possible. One, you take that and you start picking it. The seller will be silent. So you are ascertaining the goods, you are separating it, and the seller is okay with it. He is giving his consent to the separation. That is the first way. Second way, you stand still. The seller will pick up the good tomatoes for you. That is what is meaning of what? When the goods are appropriated, separated, when the bulk of goods are there, the goods that belong to you should be separated. That means appropriated. Who should appropriate it? Either the seller should appropriate it or the buyer should appropriate it. Understood this one? All of you? Done. Next one, delivery to carrier. What do you mean by delivery to carrier? Sir, at times what happens? I'll tell you my cousin runs one food brand. Yeah, they do this homemade products like the small scale industry, pickle, this papads, sambar powders, and all that. He runs that. Now, he got one order from a different place. Now, of course, I would say he has started it like it's been 2 months or something like that. Now he get an order. Now, someone messaged him that I want so and so kgs of this powder, that powder, pickle, and all that, and they have made the payment. Now, what has this person done? He has said, okay, he has gone to one of the couriers. Let us not take the names, but he has gone to one of the courier. Courier people, right? So he has gone to them. He has given the box. The box has been now delivered to the buyer. Seller has given it. My cousin has sold it. He has given it to the buyer. The buyer opened it. 2 powders, that is sambar powder and something, has opened in the transit. The boxes are opened. So when the buyer opened the total box, everything is spilled. Now the question is, who will bear the risk? The buyer sent the pictures to the seller. Now Amazon and Flipkart, very simple. It is covered under your contract. Now my cousin has zero clue that such things can even happen. He has put all that tape and all. Now tell me what will happen. Who will bear the risk? Who will bear the risk? Courier guy? Okay. Who will follow up with courier guy for compensation? Seller will follow or buyer will follow? Seller, not buyer. That's where I say, you have read this provision, read it. What does it say? When is the ownership passed? Read. Delivery to carrier. Seller, my cousin, has given it to the courier. Let us imagine some example. Say DTDC. I have given it to DTDC. When goods are delivered to the buyer or carrier or bailee, whether named by the buyer or not, meaning buyer might have not chosen it. It is a random guy. What are they telling you? Property is unconditionally appropriated. That means what? Ownership is passed. Hello, who will bear the risk? Buyer has to bear the risk. As per the law, my duty was to give you goods. Delivery risk will not be on me. Is what the law says. Again, I told you day one only. Law, what law says? Sometimes you will feel, sir, in reality, that is not how it is happening. Agreed. Because in reality, customer is the king. When law was written, customer was not the king. Today, for me to be in competition, I should still smile and say, oh, is it, sir? Okay, sir, I will bear the risk. That's how the Amazon and Mitra are able to survive. If not, there are people who are using the product and returning. No, we have to still smile and accept it, right? Yes or no? I don't have a choice. Customer is the king. To be in competition, he has to do it. But what does the law say? Law says your duty ends when you give a right product to the carrier. There ends your duty. Hello? Pakana, I only wrote this point and sent an email. Who will bear the risk? Because the cart value was what, around 1,800, 2,000. This fellow would have made profit of the entire week or something for 2,000. If it is gone, it is gone. He said, what to do? I said, see, there is one point, a section, done. But I said, for goodwill, you still say this and say that I will bear it as a goodwill. Do not do it for free of cost. At least tell, communicate, and then give it for free of cost. Now, on his website, he has this point. Any damages incurred during the transit will be completely the buyer's responsibility and not the seller's responsibility. It is there in his website today. Yes, sir. Understood? Personal branding. Okay, understood? Hello. Next one is called sale or return basis. What is my sale or return basis? All of us come here. Amazon, Flipkart. When does the ownership pass? After receiving the goods. After buyer receiving the goods, ownership will pass? Yes, sir. In my case, that is how it will pass. Who cares how it passes for them? People, sale or return basis. If you are saying ownership will pass after you get the goods, imagine if there is a hole in the shirt. What will you do? Immediately. Why? You are the owner, no?
Sir, it is different thing, sir.
That's what, you are the owner, no? You said it will pass when I receive the product. You received it, you are the owner.
You want it back and they are receiving.
See. His logic is correct. What is your name? Pramod. Pramod says, sir, when they receive it, now they will be the owner. I will send it back. They'll again give it to me. I am the owner. Huh? Yes, sir. People sale or return basis, people always remember for the ownership to pass, any of the three things should happen. What is that? The first thing is the buyer has to give the acceptance. That is in 7 days. I have 7 days time. In the third day only I say that this product is good. I will keep it. I have given my acceptance. The second one, people, there is a time period. That is 7 days is there for me to return the product. I do not return the product in 7 days. From the 8th day, it is understood that I am the owner of it. I have accepted it. The third thing, you do something equivalent to an acceptance. What do I mean by that? In third day, you will use it or you will gift it. When will you gift it? When it is yours is when you will gift it. You will not give someone else's product, right? So in these three cases, in sale or return basis, the ownership will pass. They will ask you in the exam, remember and go. In sale or return, the ownership will pass. Upon acceptance, second one, upon the reasonable period is done. The third one is you do something equivalent to an acceptance, pledge to, gift to, etc. Hello. The last one, people, reservation of right of disposal. What do you mean by reservation of right of disposal?
Seller will be rights. He still has the ownership.
Now, for example, reservation of right of disposal means people, the seller will say, see, if I give it to the carrier. Now, for example, I'm taking wrong example, but I should not take. Okay, remember. Now, I have one clothing brand. Yes, sir. Now, whenever people, ask for the goods, of course, in India we have both. Even though we have UPI payments, people will still give cash. Handling cash is very, very difficult. For example, I sell this clothing brand, I sell this clothes. If someone is paying by cash, I need to pay 5%, close to 5% overall for the delivery company for managing this cash flow. That's why nowadays, wherever you see, if you are doing cash, they will collect 50 rupees extra from you. Why? Because we have to pay. It is not something that is coming to me. The delivery companies charge it on us. Yeah. Now, what do I say? Now, say for example, there are certain people who will place exchange, meaning they might have purchased L size. You guys will get an option to do XL, meaning you can return it, you can exchange it. Now, I will tell my delivery guy clearly, a person has tried to return the L product and he wants XL now. Now, what do? I will tell my delivery guy clearly, meaning we have tied up with a delivery agent called as Shadow Fox. We clearly have an instruction. When we are selecting shipment, I get an option to click it. I will click shipping. I have to deliver it to a particular place. Now they will clearly ask me, is there any instruction to be given to the delivery guy? It will be clearly written. Now what is the instruction I will say? Do not give the product until the product that the buyer is returning meets with our return policy. What do I mean by that? The tags should not be torn. The product should not be used. Check for stains. Because I'm telling you, very, very unfortunate. Our Indians only. I'm not even kidding. People will take it for 1 or 2 day photo shoot. They will return it. Now I am only a receptor. I know. I get it back. It will be completely used. It will stink. Yeah, our Indians will do. They can do anything. Yes, ethic and all somewhere ground for it to go. So, but yes, that's how the online business survives. Now, what we have to do? We have to do a bio wash for the product again. And technically, if you ask me, it's a used product. Now you know wherever you are getting sale. I'm telling you the complete system in front of you. There are agents who will buy such returned products from us for a throwaway price. It will be taken for kgs. 1 kg will be what? 80 rupees. So in that 1 kg, you will get 4 t-shirts, 5 t-shirts. They take it from us. And that is what you guys will see in all these places where you will still have tag. You know that it is new. That's how it is done. That's the system. Understood? Yes, Now, what is reservation of right of disposal? Technically, in my previous example, my cousin's example, what did I tell you? Me giving it to a delivery agent, ownership is passed. Here, what am I telling? Ownership is not yet passed. Hey, Shadow Fox, wait. I've given you the product, but still I am only the owner. Until what point? Until there is an instruction. What is the instruction? If at all the return policies, that is the product that the person is returning, does not meet our standard, then bring back the product. Do not deliver. It's an instruction given. So I have reserved the right of disposal. I am only the owner until that particular instruction is met. This is only called as what? Reserving the right of disposal. Hello? So ownership will not pass until that particular criteria is met. Hello, clear? Done. Next one, risk transfers with ownership. This rule has following qualification. What is that? Yesterday only I told you this. If delivery has been delayed by seller or buyer, goods shall be at the risk of the party in default. Where did I give you the example? Attempted performance. Flipkart tried to deliver you the product. You were not there. The product went back. Now any damage happens to the product will be on the buyer, not on the seller. Correct? Next one. Remember, duty and liability of the seller or buyer to take care of the product as a bailee will not come to an end. What do I mean by that? Now, or take the car example. Where was the car? Have you taken enough care of the product? If you have taken enough care of the product and still this happened, then they are telling you seller has taken enough care of the product, then the seller can't do anything. Buyer will be responsible. But seller did not take enough care of the product. Macha kept it wherever he wants. Then they are telling you people, the seller has taken enough care of the product. If still something happened, then buyer. If seller has not taken enough care, seller only will be responsible. That's what is called as duty of the bailee. Now, for example, to tell you, today you place the written request. Agreed? You have clearly said, I don't want this product. Who will be the owner of that shirt today? Seller only. Now, when it is with you at your home, imagine coffee spills over it. Who will be responsible? Because it is your duty, negligence. As a bailee, you are responsible to take enough care of the product. Correct? Hello? That is what they are trying to tell you. Understanding that? Okay. Who can transfer the title? Nemodat Kwadana Beta. What do you mean by that? No one can give what they do not have. If I am not the owner, I cannot give you ownership. Yesterday only we saw. If at all A is selling B a stolen goods, B can never keep it. B has to give it back to the rightful owner because A does not have ownership. How can he give you ownership? Hello? Agreed? That is what they are telling you here. But this rule has certain exceptions. First exception is what? Mercantile agent. What do you mean mercantile agent? In the business, you appoint someone else. Now they will be taking care of the product. You will not be taking care of the business. So in a mercantile agent, nothing but in a business, the principal will not sell. Someone else will sell it on behalf of the principal. Whether will you get the ownership? Answer is yes. Example, sir, car, second-hand car showroom. You do not meet the seller. Real estate, you do not meet the seller. You meet the broker. But him selling is like seller selling only. That is what they're telling you. Hello? Next one of the joint owners. What do you mean one of the joint owners? Joint owners. Sir, there are two owners. It's called as co-ownership. Whenever there are two owners, if one of them is having the possession of the product, if that person sells the goods, it is considered as a valid sale. Technically, both of them have to sell, no? Hello? If the goods are in the possession of a person who is selling it, even if consent is not there, if consent is there, then this rule will not apply at all. Consent to keep the possession. So, A and B are the co-owners. Example, anyone is staying in PG, roommates. Any two people staying together now. Now you both are staying together. Okay. Let us imagine you guys invest in something. Let us imagine one fridge. Sir, chill. We should have fridge. Okay. Together you invest. I invested 5K, you invested 5K. Then what are you guys called as? We are called as co-owners. Now let us imagine one of the friend, after the exams are done, goes back to home. But one friend continues to stay. Now what is happening? The fridge is in the possession of one of the friend. The other friend left. Now the other friend never came back because the other friend moved on with something else there. Now this friend also came time where she has to leave. Now she's thought I'll sell everything that is there in the room. Now the question is, if she sells this fridge to a person, Say for example, Pramod wants to buy because he wanted to test the jacket. Now the question is, if Pramod is buying this fridge, whether Pramod will get the ownership or not.
Yes, sir.
Now, don't you think there are two friends who have purchased it? Both of them have to agree, but only one friend is selling it. They're telling you it is still valid. Co-owners, one person having the possession with the consent of other. You know that I am having it. And if I give it to someone else, they will get the right to ownership. Amongst you, you fight who will get the money. But for the buyer, he will get a good ownership. That is what they're telling you. Clear? Next one. Sale by person in possession under voidable contract. What is this voidable contract? I gave you an example, if you remember. What? I don't know. Jiva's case. I said, Jiva, give me your bike. Jiva said, no, sir, I'll not give. I said, hey, give. Jiva didn't come only. Yes, sir. So that is how I threatened her. Now, people, Jiva gave me his bike. I went and I sold the bike in the first floor. Is this a valid sale? Think and tell. I took the bike from Jiva. All documents properly signed. I took the document to the first floor. I am saying that this particular bike is for sale. And someone gave me money. I transferred the ownership there. Is it a valid sale? So it all depends upon voidable contract. If at all that person, Jiva, has not cancelled the contract within time, then people, the world will not know that all this is void. The world will think, yes, on the documents, I am the owner. The contract will be valid. So whoever purchased in the first floor will get ownership. If Jiva had not acted within time, he has not cancelled the contract within time, then the person who purchased the first floor will get the ownership. Hello? Understanding? See, provided contract is not cancelled. Next one, sale by person obtaining possession before passing of the property. What is this? Sale by person obtaining possession before passing of property. What do I mean by that? Sale on return basis. I purchase something on Amazon. 10 days return period is there. That means for 10 days, who is the owner? Amazon is the owner for 10 days. Provided I have not used it, I have not agreed it, I have not done something to it. For the 10 days, Amazon continues to be the owner. Agreed? Now, sir, I take this, I give this to Mr. B on 5th day only. Technically, I don't have ownership, but I'm giving it to someone else. Is B getting a good title? Answer is yes, sir. That is what they're telling you. A person who gets the possession before getting the ownership. In a sale or return basis, I first get possession. I get ownership after 1 week. In between, if I still sell it to someone, it is considered as a valid sale or a valid gift or a valid pledge. Correct? In sale or return basis only you would have seen this. Doing something equivalent to an acceptance. Hello? Next one. Sale by person who has already sold the goods but continues in possession. What do you mean by that? For example, people, I showed you the phone. Now, Jiva's phone. Allah. Nitish's phone. Okay, imagine like this. So for example, I'll say, people, this phone is for sale. No defects. This phone is for sale. Yes, hey, forget that. No defects. This phone is for sale. Now, people, someone said, sir, I want to buy. I said, say 5,000. He said, yes, sir, I'm okay. But I will give you after 1 week because I need to transfer the data. He said, okay, sir, I don't mind. Yes, you tell me, is the ownership passed or not? Again, I'll repeat. This phone is for sale. How much? 5,000 rupees. I said, I'll give you the product after 1 week. He said, okay, sir. But do you want to buy? He said, yes, sir, I want to buy. I'm interested. Yes, I want to buy. Now I'm asking you, is the ownership transferred or not? If the answer is yes, the ownership is transferred. On what grounds you are saying it is transferred? He has said yes, Sante. On that ground, ownership is transferred. Provision. Ownership is transferred or not? No. Why not? No. I mean, why no? It's not in deliverable state. So according to you, what do you mean by deliverable state?
The deadline inform that it is done, then it will be transferred.
Okay, I will tell now. Nitish, the data is transferred. Come and pick up the phone. Nitish says, sir, today and tomorrow I'm not feeling well, sir. I'll come to class on Monday. I'll pick it on Monday. Is the ownership phone is still with me? Is ownership transferred? Possession is with me only. Ownership is transferred. Now, people, what I will do? Nitish said I will collect the phone on Monday. Correct? Now again I gave it a try. People, this phone is for sale. Anyone wants to buy? Pramod comes and says, yes, sir, I am interested. Because that day Pramod did not come to class. Pramod said, I am interested. I said, how much you will pay, Pramod? Pramod said, I will pay 10K. I said, it is wonderful. If I give it to Nitish, I should have sold it for 5K. The product is still with me. Goods which are in deliverable state, ownership transferred when the contract of sale is made. Product delivered, price paid is irrelevant. Macha, car example now. When you know the phone is existing right in front of your eyes and the condition is done, goods are put in deliverable state, ownership passes, that's all. Do not think it in your real life scenario. Real life is different. Real life, we are so attached. The phone is given is when ownership is passed. No. Come out of that. If not, Hogala chapter olagada. Hello. Hitting the point. So in this case, is the ownership passed? Answer is yes. Technically, what does the law assume? The goods are in deliverable state, but the possession is with me. Hello? Now for the next buyer, I will say, I will convince him, okay, you take it for 10,000. What do I think? I will think, hey, it's okay. Nitish, I'll give 1,000. I'll tell him to keep quiet. He'll keep quiet. I will take 10,000. I'm still at a benefit of another 4,000 rupees. It's a win-win. Now, can I make this sale? Now, imagine Pramod purchased it from me. Now, my question is, who gets the ownership? Nitish or Pramod? The law is telling people Pramod will get it because people, the initial ownership, the documentation, everything still says I'm the owner. The product is also will be with me. It's very difficult for the second buyer to make it out that the contract of sale was already made. How will Pramod find it out? Every place it is my name written. How will even Pramod get to know this? Caveat emptor, okay, how will he find? How will he identify? So that's why the law is telling you, I will protect you. See here, that's what they are telling you. Try to read. Sale by person, me, who has already sold to Nitish, but continues in possession. I still have it. And I sell this to someone who, Pramod, buyer acted in good faith. Pramod does not know all of this happened. The buyer will get a good title. Pramod will get a good title. Now, what is Nitish rights? That is not given here. But what can Nitish do? Nitish can file a case on me. Breach of contract. Hello. Sir, this is too unfair, sir. It is unfair. That point is coming under exception. It's not a generic rule. I'm not telling generally this is how it is. It's an exception. We have to protect Pramod also, no? Hello. Next one, estoppel. What do you mean estoppel? Phone. Nitish phone. I told no, I sold. Can Nitish come and stop me? I'm the owner. Yesterday's case, I took Nitish's phone. I sold it to you. Someone purchased it. I don't know. I said, come and collect it after the class. Nitish stayed quiet throughout the conversation. Nitish has to continue to stay quiet. He can't stop me. Am I the owner? But I sold it, no. Valid, Unpaid seller. Next topic we'll do. Other acts. Under other acts also, even if a seller is not selling, someone else is selling, it is still considered as valid itself. When if it is sold by a liquidator, what is liquidator? Vijay Mallya, how much money did you recover? 14,000 crore. But Macha did not come to India in the last 13 years. How did you sell? Hey, if you have got money, someone should have sold, Noda. Who sold? Vijay Mallya is the owner. He's building UB City. He's the owner. Who sold? Someone should have sold. He did not sign even one document, it seems. How? Law has given a right. Macha, insolvent. If you become an insolvent, if you become a fugitive economic offender, Vijay Mallya Anna, what is a fugitive economic offender? A person who has to pay us money but has ran away. We give a special tag to them. We call them as fugitive economic offenders. Fugitive means a person who has ran away. Economic means money. Offender means not paid. Hello. Now our Indian courts has a right to sell the products. They sold. They recovered the money. Now someone has purchased UB City. Did they get the ownership or not? The question is, did Vijay Mallya sell it? Exception? Hello? Finder of lost goods. Whoever finds it is the next owner. Agreed? Third one is sale by pledgee. We saw bailment. If you do not repay the loan, the Muthoot, what will they do? They have your gold. What will they do? They will sell it. They'll give you a notice. They will sell it. If they are getting shortfall, they will ask from you. If they're getting surplus, they will give it to you. Hello. Last one, sir, rules regarding delivery. Buyer to apply for delivery. Yesterday only I told you, by default, seller will not deliver it to your place. Seller is bound to give the product wherever the sale is made. So if you go and buy something, say for example in that corner shop, the coffee shop, if you buy a sandwich there, where will he deliver it? He'll deliver it in ArivuPro. Why? You tell him, deliver it here. By default, it is delivered in that place unless and until a request is made. Hello? Seller is not bound to perform until buyer applies. I will deliver it there only. Hello? Place of delivery. Where will we deliver? Where will we deliver? So you guys should have been in normal class. Ragging what? No one can rag you more than what I can rag you. Come to regular class. Okay. Yes, sir. Rag andre I'll make you cry only. Okay, now see here. Illa kano sumne ಹೇಳಿದೆ. Yes, sir. Now see here. ಏನ್ ಹೇಳ್ತಿದ್ದೆ? Place of delivery. Where should I deliver? First one, macha, as per contract. Amazon, where should he deliver? I will clearly give, sir, address. Landmark, sir, but Anna will be standing like this. Deliver there. Correct? So I'm clearly telling where to deliver. As per the contract, they will deliver. Sir, what if there is nothing agreed? Where should I deliver? Example, sir. Kisan company went and entered into an agreement with the farmer. We want ಆಯ್ತು ಆಗ್ಲಿ ಬಿಡೋ ಬಿಟ್ಬಿಡೋ ಲಾಸ್ಟ್ ಡೇ ಬಿಡೋ ಎಷ್ಟು ಫೋನ್ಸ್ put it on silent mode. Okay, now people imagine Kisan company went and purchased tomatoes from farmer. Where should the farmer deliver the product? Where? There anta illi tab. Where should they deliver? First one, my question is, did you guys agree something? No, we just agreed that yes, I want to buy this tomatoes. Now what should I assume it as? Farmer will come and deliver it to me in my factory? If nothing is agreed, people, the product will be delivered. If it is a specific and existing goods, when the contract was made, wherever the product is at the time of the contract, meaning when we both entered into a contract, at that time where the product is, in my godown, it will be delivered in godown. In a shop, it will be delivered in a shop. If nothing is agreed. Sir, what if it is future goods? It will be delivered in a place wherever it will be manufactured, produced or grown. So if the parties are silent, then they are telling you the product will be delivered in the land wherever it is grown. If it is silent, understood? If contract is made, as per the contract. If nothing is made, wherever the products are or wherever the products will be manufactured. Example,
I enter into a contract to make a sofa with a carpenter. If nothing is agreed, or if it is agreed, generally agreed, where I will have to go and get it delivered at my home. If nothing is agreed, I'll have to go to his warehouse, wherever the carpentry work is made. I'm supposed to collect it there if nothing is agreed. Hello? Next one, time of delivery. Time of delivery, always within reasonable time. First, go as per your contract. Amazon says, I will deliver it to you within 3 days. Deliver as per the contract. Nothing is agreed. Deliver within reasonable time. Hello? Next one. Time for tender of delivery. What do you mean by time for tender of delivery? Tender of delivery means, people, the seller asking the buyer, can you please deliver the product? Tender for delivery means, people, seller asking the buyer, can you please deliver the product? Can such request be entertained by the buyer? Can it be entertained? I mean, by the seller. What did I say? Can buyer making a request to deliver the product to the seller? Tender for delivery means buyer making a request to the seller asking, can you please deliver the product to my place? Now, is seller liable to this request? It is, I'm not liable. I might take it up. It is my discretion. But remember, seller need not have to deliver the product if the delivery instructions are unreasonable. What do we mean by that? Can you please deliver the product by tomorrow morning? I want it today. By today evening, I want it. If the request is unreasonable, the seller can reject that request. That's what they're telling you. Such demand will be treated as ineffectual unless asked in reasonable time. If the buyer gives me crazy deadlines, I'm not supposed to take up that contract at all. I'm not bound by it. Hello? Okay. Next one. Goods in possession of third party. We already saw this. Constructive delivery. How will the delivery happen? Acknowledgement. If you remember. Hello? Installment deliveries. Remember, by default, the buyer is not, what is that? The buyer is not under an obligation to accept the goods in installments. For example, if I buy a car, one will come today, next will comes tomorrow. I'm not allowed to take the goods in installments unless agreed by the parties. If parties are okay, it's okay. But by default, I'm always expecting the whole contract to be delivered at once, not in installments. Next one, delivery to carrier is considered as delivery to buyer. I told you my cousin's food thing. Deterioration during transit. Yesterday only I told you. Who bears the risk? Deterioration during transit. If it is a mistake of the seller, it will always be on the seller. If it is a mistake of the buyer, it will be on the buyer. But sir, if both of them are correct, in Indian Contract Act we saw, it will always be on the carrier. Yesterday we saw the Apple case. If at all I delivered the apple today, I can sell the apple at 300 rupees. You delivered the apple after 5 days. There is a value deteriorated. Who will bear it? The carrier has to bear it. Hello. But sir, it so happens at times that whenever some products are purchased, the products are purchased from a distant place, meaning far. Now it is common sense that there will be a deterioration involved. It is a common sense. For example, whenever you guys order ice cream on Zomato or Swiggy, anyone orders? You order? Yes. Now imagine you ordered ice cream, but milkshake came. Is it okay? Because it will melt. It will come always like that. At least once have you tried to raise a ticket? No? Why don't you try? No, wait. That ice packet will be given to you only when the seller sells it that way. Meaning that gel. That is not given to you by Zomato or Swiggy. It's the ice cream wala. That means you are buying it from a premium place. Buy Cornetto or whatever your Magnum on Swiggy, Blinkit or something, Instamart. Now you see whether you get that gel. You will not get it. They try their best. Of course, they are trying up with whatever equipment, the bike, the foil, they are trying their best. Nowadays, they carry one special pouch to keep these items. No matter what said and done. Now you tell me, you order an ice cream, it is melted. Can you guys file a ticket on the Swiggy or Zomato? Ask for money back. Will you get it? Why? Hey, you purchased ice cream, da milkshake came, huh? What you guys? Huh? So remember, people, you cannot fight a case. Why? Deterioration during transit. Common sense. Ice cream will melt. Even then, if you are buying it, it is the risk of the buyer. Seller can't do anything in this case. Hello? Understood? Pakka na? So for example, whenever there is import and exports involved of iron, ship route, ship, if they're selling something by ship, on a bare minimum, ship takes around 40 to 50 days to reach your destinations. Bare minimum of 40 to 50 days. Imagine iron, you're selling iron bars. You shipping it in a sea route. It going for 40, 50 days. Don't you think iron will definitely have rust involved? That too, you're traveling in a sea route. The moisture will be there. The content, salt content in the air will be there. There will be rust involved. Now the buyer opened. He has ordered for iron. When I sold, it was perfect. But when you open it, there will be rust. Can I cancel the contract? That is what is this? What is this condition you are seeing? Deterioration during transit. See what do they say? Goods deliverable at a deterioration incidental. What is by incidental? Ice cream will melt. It's common sense. Incidental means the product's nature is that if you still order, then the risk is on. Understood? Hello? Buyer's right to examine the goods. Flipkart, Amazon, that open box delivery. I have to give my OTP and we give it with checking. Correct? Buyer if not already examined. Did I check the phone? So he has to give me an opportunity to check the phone. I checked it also. Has to examine the goods before accepting delivery. Macha, once I check it, done. Correct? Hello? Okay, last topic, we'll finish it off and go for break. Unpaid seller. Who is an unpaid seller? A person who has sold the goods. A has sold the goods to B. The product value is 10,000 rupees. B has paid 9,999. B has not paid 1 rupee. The question is A an unpaid seller? 1 rupee is not paid. Is A an unpaid seller? 1 rupee. Even for 1 rupee. The words used, people, are I will be considered as an unpaid seller if whole of the price is not paid. Whole means what? Full. Until 10K is paid, people, I will be considered as what? Unpaid seller. Agreed? Yes, all of you. So that is what they are trying to tell you. Whenever a person has given the buyer a time period to make some payment, if you do not make the payment within that time, my right will be something called as an unpaid seller. Unpaid seller will have 2 rights. One is against the products that I have, against the buyer for not paying on time. So on products, you will further have 3 rights. What is that? The first one is called right to lien. Second one is called right to stoppage in transit. The third one is called right to resale. What do you mean by right to lien? Whenever the ownership is passed, but I have told you, for example, I give you some time. Say, for example, I'll tell you, see, this phone is sold. Now, Nitish has purchased it. So, Nitish said, sir, give me time till evening. Now, first I asked Nitish, 10K, okay. Nitish said, okay, sir, 10K, I'm okay with it. Data, everything is done. Now, goods are in deliverable state. It is here. Nitish, take and go. Nitish said, sir, give me time till today, end of the day, that is today night, I'll come and make the payment. I said, okay, Nitish. Goods are in what state? Deliverable state. Have I received money? No. Is the ownership passed?
Yes, sir.
Answer is yes. Now people, 5 hours done, Nitish did not come. 8 hours done, Nitish did not come. Night, Nitish did not come. Now, by the next day, what am I called? The next day I am called as unpaid seller. Now Nitish is coming and asking, Nitish sent his friend, Macha, go get the phone, we will transfer the money. I said, Nitish, simple. Pay the money, take the phone. It is simple, concept is simple. Yes, ownership is with you, but pay the money, take the phone. Until the money is paid, will I give the product? Until the money is paid, will I give the product? Me holding the goods with me like this until the money is paid is called as what? Right to lien. The goods were with me. I retain it with me. The words, again remember, in exam you need to write these words. That is the key word. The goods were with me. I need to retain it with me until the money is paid. This right is called as people. Right to lien. Yes? Hello? Pakka? Now, what do you mean by right to lien? Right to lien is nothing but keeping the product with you until the money is paid is called as what? Right to lien. The next right the seller has people, something called as right to stoppage in transit. What do you mean by stoppage in transit? Now, for example, I told you, right? Let us imagine I sold certain cloth to a person called B through that, say, for example, through Shadow Fox. They will take 4 days or 5 days to deliver. Now, on third day, people, I got to know that B has become insolvent. But I've already given the goods to Shadow Fox. Now, they have picked it from my location. Now, they are on the way. It is not yet delivered. I will call Shadow Fox person and say, hey, B has become insolvent. Don't go his home. Come back with the product. Come and give it back to me. Now, what do you mean by right to stoppage in transit? Transit means what, people? The goods were with me, but it went away from me. Now it is with the delivery agent. But still my money is not paid. I got to know that he cannot pay the money also. In that case, what will I do? I'll call the delivery guy. I'll tell him, Macha, bring back the product and give it back to me. Remember, right to stoppage in transit can be exercised only when the buyer becomes insolvent, no other grounds. So people, right to stoppage in transit means people, right to regain the possession. I had it with me. Now I'm again telling him to bring it back. Regain and retain until the price is paid. Regain, retain. Again keep it with you until the price is paid. It's called as what, people? Right to stoppage in transit. Now, sir, I got back the goods. I wait for Nitish for until today. Tomorrow, day after tomorrow, Nitish did not pay. But as per law, I have transferred him the ownership. How long shall I wait? Law says, Macha, wait for a reasonable time. He did not come. Inform him. Nitish, today is the last day. If you do not come, I'm further going to sell it to someone else. You have notice till today. If you do not pay, then I'm going to sell it to someone else. Nitish does not come even by today, people. I have a right to resell the goods. The third right to resale. Hello. Who is the owner? Nitish is the owner because remember I told you goods which were in deliverable state. Ownership passed to Nitin. Now you tell me, do I have a right to resell it? Technically, he is the owner. How can I sell it then? Exception to Nemodat Quad non-unpaid. That is where they have written, people, right to resale by a unpaid seller. I still have a right. I can sell it. Understood? Hello. Okay. Taka seat of right to lien. What does it say? It's meaning the right to retain the possession until the price is paid. It can be exercised only when goods is not sold on credit. Or if sold on credit, the term has expired. Macha, come and give it to me by tonight. Buyer became insolvent. So in these three cases, I can always exercise right to leave. Right to sit the only last one.
They can ask you difference-based question, remember and go. Hello. Termination of lien. When does lien come to an end? First one, delivery of goods to the carrier or bailee. Correct? Huh? I had it with me. I give it to Shadow Fox. Lien comes to an end. Done. Buyer or his agent obtains the possession. I have given it off to Nitish. That's all done. Where is right to lien? Third one, seller waived the right of lien. I said, okay, Goda. Nothing but people give up. Fourth one, people estoppel. Estoppel means what people? By conduct. I said, Nitish, I'll keep it here. Come make the payment and take it. But Nitish was about to take it. I did not stop him. So, waiver and estoppel are one and the same. Waiver is express. Estoppel is by conduct. I keep quiet. That's all. So, by this, effect of lien will come to an end. Hello? Okay, next one is transit. What is stoppage in transit? Whenever the goods are in the transit, I have a right to regain the possession. It can be exercised only. Stop the goods while in transit and you will regain the possession. And you will retain it until the price is paid. Correct? When does the transit come to an end? When the buyer or bailee obtains the delivery. That means people, once the goods are given, even the transit will also come to an end. Of course, right? Hello. Next one, carrier or bailee acknowledges to the buyer that he holds the goods for him and seller has not reserved the right of disposal. What do you mean by this? The acknowledgement. Nothing but the constructive delivery. The third party said, sir, the goods are reached or I am holding it for you. When that call is made, they are telling you people the delivery is completed. The right of stoppage in transit will come to an end. Sir, what do I mean by that? Let us imagine the A to B. A is sending some goods to B. You can send it no on Rapido. You can send parcels, right? So I call a Rapido guy. He comes near my home. He picks up the parcel. Once he has crossed halfway, he has almost come near the B's place. Now Rapido guy has come here. Whom will he call? A or B? Whom will he call? You will clearly be writing the name, recipient's number. He will call and say, sir, I have arrived. They're telling you delivery is complete. Acknowledgement. Technically, where is the goods? The goods is in the possession of the third party. That is a Dunzo or a Rapido. Correct? It is neither with me nor with him. Now, technically, you tell me who is having the possession. Is it the seller or the buyer? It depends upon the acknowledgement. The moment he called and said, sir, I have arrived. Your products have reached. It is technically not in my hand. But I'm telling you, the delivery is completed. Rapido will not listen to A now. He will listen to B only. Is what they're telling you. Understood? Hello? Okay. Next one, goods delivered to the carrier hired by the buyer. This is the simplest one. The buyer only sent you the delivery agent. He will of course listen to him. We do not have any control. The transit will come to an end. Carrier wrongfully refuses to deliver the goods to the buyer. What do you mean by this wrongfully delivered? I mean, wrongfully refuses to deliver the goods. Wrongfully refuses to deliver the goods. Now, for example, people, has it ever happened to you? You are at home, you do not get a call, but you get a message from Amazon or Flipkart, attempt to do delivery failed. Have you ever got it? That is only called as what people wrongful delivery, wrongful refusal of delivery of goods. You were there. You had a right to pick it up. The delivery guy wrongfully refuses to deliver. Your mistake itself is not there. You were not even contacted. Technically, you have a right to receive it. But the delivery guy refused to deliver. Why? Because of whatever reason, he has refused to deliver. Now, in that case, they're telling you, transit comes to an end. Meaning what? Amazon guy has sent you a message that we attempted the delivery and the goods are taken back.
Technically, if you think the goods are still with the delivery guy, it is still in transit. The seller can call it back. But how is he having the goods in transit? They're telling you by mistake. It's not rightfully, it is wrongfully. They're telling you transit comes to an end. Amazon can no longer recall the goods, is what they're telling you. Understood all of you? Hello. Okay. Part delivery considered as full delivery. For remaining goods, the transit comes to an end. What are those people? Okay, you can imagine like this people. Part delivery. Let us imagine I'm selling 1 lakh kgs of tomatoes. 50,000 kgs of tomatoes are delivered. Another 50,000 kgs of tomatoes are on the way. They're telling you for the first 50,000 kgs, the right to transit has come to an end. But for the rest of the 50,000 kgs, whichever is on the way, for that you can exercise right to stoppage in transit. Part delivery means what? Have agreed to deliver a huge quantity. In that, I have delivered only the part of it. Rest of it is on the way. Whatever is delivered, I cannot recall it. Whatever is on the way, I can stop it. Agreed? Yes or no? Next one, goods delivered to the ship were charted by the buyer. This generally happens, people, in the case of export and import. Same as this point. This we are taking a simple roadway. This we are taking it in the import and export. Imagine you have given it to the shipper. The ship was not hired by you. It was hired by the buyer. In that case, people, the goods are agreed to be delivered to the buyer. Agreed? For example, I'm saying when we are also making sale, there are a couple of buyers in a different country. There are two ways to handle it. One, I go and I do the complete export part. Second one, the buyer in the country will tell me, you have to give the consignment to this place by this time. From there, they will take it. Both the types of sale will exist. Yeah. Now we fallen. I don't know any ship or any agent. So what will I do? I go to a person, I deliver it there. From there, the buyer will take care of it. I get the point, all of you. That is what is goods delivered to the ship charted by the buyer. How stoppage and transit is affected? You personally go and get back the goods, or you call them to bring back the goods. Both are valid. Effect of subsale or pledge by the buyer. What do you mean by subsale? Sir, A has sold the goods to B. B has sold the goods to C. B has not made the payment, but C has made the payment. Now the question is, should A give the goods to C, or whatever my rights as unpaid seller are, that is lien or stoppage in transit or right to resale, what will happen to those rights? Will it come to an end? Now this only is called as what people subsale. I have agreed to sell it to you. I have agreed to sell it to Nitish. I have not yet given the phone. What has Nitish done? Nitish has gone and sold it to someone else. Macha, there is one phone, so and so model. I will sell it to you for 15,000. So Nitish has agreed to C. C has given money to Nitish. But Nitish has not given money to me. My question is, what is my right? Can I still keep the goods with me? C is coming and asking the goods from me. Sir, Nitish said your phone is for sale. I made the payment also. Can you please give me your phone? The question is, should I give my phone to Nitish? I mean to C. Am I under a liability? So remember people, by default, subsale is not valid. Meaning my right of unpaid seller will not come to an end. I will tell C, please come back. You go and question Nitish. You have nothing to do with me. My rights of unpaid seller will not come to an end. Unless, let us imagine, Nitish purchased the phone with me this way. I said, people, anyone wants phone? Nitish said, sir, yes, I want. I said 5,000. Nitish said, sir, do one thing. I will further sell it to someone else. I will get the money and then I will pay you. I said, okay, Nitish, I don't mind. That means what? I have given my consent for subsale. I have agreed. Now, if C has paid money to B, B has not paid money to me. It is still okay. I can't do anything. If C comes and asks the goods from me, I have to give because I have agreed for subsale. If I have not agreed, then people are not under a liability to give it. If I have agreed, I have to give it. Hello? This is only called as effect of subsale. Clear? Pakka? Okay. The next one is effect of pledge by buyer. Now, what do you mean by this? Pledge or sale. Try to read this, see if you guys are understanding something. A document of title. Read that. People, there's a go down. The go down full has clothes. Full go down is full of clothes. A sold the goods to B. The go down has the go down certificate. We call it as warehouse certificate. Now B has not yet paid money to A, but A has given this warehouse certificate, the go down certificate. I've given it off to B. Now, what is this document? What is this certificate? Remember, people, it is a document of title. Whoever goes and gives this document, people, you will get the ownership. You will get the goods. Agreed? Hello. Now, people, in this case, what will happen? Now, he will go and give the goods to the go down. Go down person doesn't care whether what if the money is paid or not. We do not care. Now, people, that is what they're telling you. If at all the document of title is passed to B and B has given it to C. Now, how has B given it to C? He might have given it in two ways. One, he might have given it as a sale. Second one, he might have given it as a pledge. Meaning B has taken loan from C based upon this clothes. I have given it to B. B has taken loan from C, keeping this as security. Can happen, no? I hope you are understanding illa. A has given the goods to B. Now B has further done a subsale, or B has taken loan from C by giving something as security. What has he given? He has given this stock as security. Hello? Now, sir, B has not paid me money. What is my right? In a document of title, if we have given it to B, B has also further given it to C as a sale. Your right of unpaid seller comes to an end. Full stop. Sir, A has given document of title to B, but B has not sold it to C, but just to pledge it with C. As a security I've given. What have I given? I've given this document as a security, and based on that I've taken loan. Now what A can do? A can just go and request C. Sir, this person B has to give me also money. I understand he has not given you also money. But sir, if you have any other property of B with you, can you please first sell that and recover your money? And if it is still pending, some money is still there, then you please take it from my goods. But if the other earlier goods only can repay your money, can you please give this goods back to me? Because even my money is not paid. You can just go and request. They can ask you this whole scenario. That is what is this? In a sale, the lien or stoppage in transit is defeated if you have given document of title. But if it is a pledge, the lien or stoppage in transit may be exercised by. It's a request. It's not a demand. It's not your right. I hope you're getting that. Done. The last one, sir, right to resale. Sir, I've got back the goods. What will I do with the goods, people? Remember, people, the goods can be of two types: perishable, non-perishable. Imagine apple phone. Apple is, I'm saying, okay, orange. Orange and phone example. Orange is a perishable goods. Now, if at all it's a perishable goods, I need not even tell the buyer, Macha, if you don't come and repay, I will resell it. Because for me, every day matters. The orange prices will keep on decreasing. I need not even ask the first buyer. I can directly go and resell the goods without even informing them. But sir, in the phone case, goods are not perishable. I can wait for some time. The law expects me to inform Nitish once before I sell it to someone. Give him a final notice. I give you last 2 days. If you do not pay, I will give it to someone else. Please inform. Sir, now 2 scenarios. I informed, I did not inform. I informed, I did not inform. If I did not inform, now I sold this phone for 5,000 rupees with Nitish. Now I did not inform. I again came back to the class. I auctioned it again. You guys thought, oh, 5,000 it did not go. Now you guys auctioned it for 3,000. Technically, the product went for a lower price. Now, people, I will file a breach of contract with Nitin, ordinary damages. I will ask Nitish to pay me 2,000 rupees. If I tell Nitish, if I've given him a notice, I have a right to recover the loss. Sir, what if I did not give notice? I cannot recover the loss. Sir, what if, imagine I did not tell Nitish I'm selling the phone. I came back to the class. I'm again telling people this phone is for sale. Now it went for 10,000. But I did not give notice to Nitish that I'm selling it. I sold it for a profit. The profit, I cannot keep it. The profit should be given back to Nitish. They can ask you what is the effect of resale. What happens at the time of loss? What happens at the time of profit? When the notice is given, when the notice is not given. Important, remember and go. Hello? Pakana. Sir, perishable goods. Should I give notice? Whether you give notice or not, whatever is the loss, you can definitely recover. Which one? In the case of perishable goods. In the case of perishable goods, whether notice is given or not, it is the same effect as if in this case, whatever we have given here. Meaning, whatever is the loss, I can recover. Whatever is the profit, I can retain. It is assumed that it takes the effect of notice is given. Sir, when else notice is not required? In the contract only I have clearly written. If you do not give it to me by this day, I will automatically resell it. That time also, I need not give the notice. Any loss, I can recover it. Any profit, I can keep it. Clear? Hello? Done. Last one, right against the buyer. What is the right I have? I can file a suit for price, meaning I can file Nitish, give me 5,000 da. Damages, Nitish, give me 2,000 da. Correct? Next one, I mean, of course, all the other damages, whatever we have seen in Indian Contract Act, special law, exemplary, nominal law, as the case may be. Hello? Next one, repudiation of contractor. Nitish, if you come tomorrow, you will not get it. I'm cancelling the contract. Today is the last day. Last one, suit for interest. I've paid people 5,000 rupees. If Nitish has given today versus Nitish gives me after 1 month, are they both same? Income tax, sir. I told you yesterday. You had given in 2014. The fine would have been, say, 97 lakhs. You're paying tax today. Then pay with interest. Hello? Agreed? So even I have a right to recover it interest. Hello? It's the last one. Suit for interest. Agreed? Next one. Right of buyer. What is right of buyer, sir? Now, when a seller has some rights, even the buyer also has certain rights. What is that? Damages for non-delivery. Meaning, if I take the money, but I did not deliver the product, he can also file a case on me. Suit for specific performance, which I have already told. Antique items, goods of some special importance. I can say, as a buyer, I don't want money as compensation. I want goods only. That can happen only when the goods are of some special importance and money is not a valid compensation. Only then they will order specific performance, not generally. Next one, sir, suit for breach of warranty, nothing but claim compensation. That can be done. Repudiation before due date, he can also cancel. Last one, suit for interest. Sir, I have paid advance of 50,000. You are giving back the 50,000 today. 1 month you kept it. Give me interest on it. He can ask in return. The last one is called as auction sale. What is auction sale? Auction sale is nothing but the goods sold in a bid for a highest price. It's called as an auction. Yes or no? The auction can be always, remember, the goods can be sold individually or in lots. Meaning I can sell one by one product. I can combine every product and sell. Anyways is allowed. Completion of sale. What is completion of sale? In auction, when is the sale complete? It depends. It depends upon the tradition the auction house is following. It can be hammer, it can be bell. Everyone follows their own thing. 3 times hammer is considered as sale. It's a hammer tradition. Few people will follow bell. It can be as the case may be. The next one is right to bid may be reserved. What do you mean by right to bid may be reserved? At times the seller itself can reserve the right to bid. It generally happens. I'll give you an example. There is say imagine A wants to sell all his goods. So I went and I contacted an auction house. Auction house is like people and agent. Yeah. Now they know the value of each item. Now A said, can you please sell all my goods on an auction? Now the auction house agreed. The people on the day of the auction house feels that A has one product, which one, let us imagine an antique clock. The auction house feels this is a really good product. They only want it. Can they keep it? Are you getting my question? Auction house who has done this business for auction for 10-15 years, they know the value of the clock. Can they only keep the clock? Can they do it? Remember, if they want to do it, they have to reserve the right to bid. The auction house has to intimate the entire public or have given the notice. No, in that I should be telling one representative from my company will also participate in the bid. This is only called as right to reserving the bid. It can be that. It can be this. Majority cases will happen this way. Understood? Hello? Now, can they participate? Yes. If they think value is good, they will participate. Why not? Can't they do? Why? They are disclosing and participating. That's why. If I do not disclose, then what will happen? Now it is called as what? Voidable. If the buyer gets to know, if a person has participated without telling, then I can consider it as a voidable. I can consider the entire contract as void. I can ask back for money. Getting the point? Hello? Next one. See, if notified, it's legal. If not notified, agreed? Yes, sir. Reserved price, base price from which auction starts. People, there are too many types of auctions, people. One is called as closed house auction, open house auction. You know what is by closed house auction? Closed house auction means you cannot participate in the auction without an invite. Random public cannot participate. Open house auction, anyone can come and participate. There are many types of auctions. Understood? Okay. If it is a closed house auction, a person comes and bids it without a right. The sale is invalid. Yes or no? Why am I telling this people? Exam question. I'll show it to you. We'll see that question. Pretended bidding. What do you mean pretended bidding? CSK does not want someone. Say for example, they don't want the Jadeja. Who is Jadeja? Where is he now? Oh, that Farm Noda. Huh? Oh, Sanju Samson is back. Okay. So much happened, Okay. Now, people, now CSK does not want Jadeja. But in the auction, they do not want to give it away for a less price. What will they do? Now RR wants Jadeja. They said we will buy for 5 crore. CSK, we don't want it, but still we'll say 8 crore. RR wants it, they'll say 10 crore. We don't want it, we'll still say 12 crore. We will take and keep it in a place where we'll say, okay, now take. This is called as what? Pretended bidding. If I can prove someone did pretended bidding, that contract will be voidable. Meaning, I can say, come back, do the auction from the scratch. Hello. Pakana. Okay. Go for a break income. Yes, people. Okay, let us see some questions and then take up, we'll continue the class. Till where had we done that? Any idea? Bottle and all was done. M Limited was done. M Limited contract with Shanti Trade done. Okay, done. Sheena. Sheena, you know Sheena? No, you don't know her? Okay, then. Sheena was a classical dancer. She entered into an agreement with Sheetal Vidya Mandir for 60 dance performances. As per the contract, she was supposed to perform every weekend and she will be paid 10,000 rupees per performance. However, after a month, she was absent without informing due to her personal reasons. Answer the following questions as per Indian Contract Act. Whether the management of Sheetal Vidya Mandir have the right to terminate the contract?
Yes.
Do they have? Yes, they have. Because it's a breach of contract? Yes or no? If the management of Sheetal Vidya Mandir informed Sheila about its continuance, can the management still resign the contract after a month on this ground? Subsequently, if the management of Sheetal Vidya Mandir informed Sheena about its continuance, can the management still resign the contract after a month on the ground? Subsequently, possible? Yes or no? So remember, people, once same like misrepresentation. You had a right. If the person did not come on time, if the person did not come for the performance, you have a right to cancel. Cancel it and go ahead. You did not cancel, you gave her a chance to continue on the same ground. Again, subsequently, you do not get a right to cancel. Hello? Can the Sheetal Vidya Mandir claim damages that it has suffered because of breach in the case, in the above case? Possible? Can they claim damages?
No.
Can they claim or not? See, yesterday I told you, no? You got to know the vibe. You guys understood what I was talking about? Vibe. Vibe. Understood? The answer, can I claim compensation?
Sir, I think no, sir, no, sir, no damages.
Huh? No damages? Breach of contract, whether you suffer damages or not, can I claim compensation? Answer is yes, I can claim compensation. No? Yes or no? Breach of contract, whether you suffered damages or not, end of the day, it is a breach of contract. Ordinary to nominal, whatever it is damage, yes, you can claim compensation. Why can't you claim compensation? Pramodo, as part of such a Sheetal client can suffer because in light of the provision of Indian Contract Act 1872, answer the following. A and B now. A and B entered into a contract to supply a unique item, the alternate of which is not available in the market. A refused to supply the agreed upon unique item to B. What directions could be given by the court for the breach of such a contract? Suit for specific performance. It will still come under breach of contract. Remedies, I can seek specific performance. Antique item, unique items. This is what I was talking about. Hello. Mr. Murthy was traveling to Manali with his wife by bus of Himalaya Travels Private Limited. Due to some technical default in the bus, the driver has to stop the bus in a midway in cold night. Driver advised the passenger to get the shelter in nearest hotel, which was at a distance of only 1 kilometer from that place. The wife of Mr. Murthy caught cold and fell ill due to being asked to get down, and she had to walk in the cold night to reach hotel. Mr. Murthy filed a suit against Himalaya Travels Private Limited for damages for the personal inconvenience, hotel charges, medical treatment for his wife. Explain whether Mr. Murthy would get compensation for which he filed the suit.
No, no,
Yes or no? Sabas. No. Why?
Sir, you can only get the claims for ordinary damage, not extraordinary damage like the health issues and medical treatment.
Medical treatment, I cannot get it.
Yes, sir. Sir, you can get, sir.
Uh-huh.
There's a damage for non-graduate students, so they will get
They'll get
expenses.
medical expenses also.
Yes, sir.
Medical expenses also will get. Pramod?
Yes, sir.
Sir, if I was there, I will give. Correct, Pramod?
I will get, sir.
I will get, sir. Whether they will give or not, I will get. People remembered. Now, my question, imagine that if 40 people got down, 40 people walked from that place to that place. Did everyone got cold? Or only this wife got cold? Extraordinary case. That means what? Special damage. Remember, by default, you will never get special damage. Special damages will only be given if at all there was any intimation given. Nothing is given here. Now, because there was a breakdown, did everyone take shelter in hotel? Answer is yes. Why did we go to hotel? Because the bus did not work. Now, the health issue was somewhere which you could not foresee. So, hotel directly related. What else they have given? Personal inconvenience, hotel charges. Yes, it is directly related. Everyone personal inconvenience. But people, medical treatment, you are one of a case. It's not ordinary. It is special. So what will you get? You will get what is directly related. Hence, in the given case, Mr. Murthy will not succeed in his claim. Mr. Murthy can claim only ordinary damages, which was directly related and proportionate to the damages caused. So hotel, yes. Medical, no. Clear? Huh? Hello. Mr. Y, age 21 years, lost his mental balance. After the death of his parents in an accident, he was left with his grandmother, aged 85, incapable of walking and dependent upon him. Mr. M, their neighbor, out of pity, started supplying food and other necessaries to both of them. Mr. Y and his grandmother used to live in the house built by his parents. Mr. M also provided the grandmother some financial assistance for her emergency medical treatment. After supplying necessaries to Mr. Y for 4 years, Mr. M approached the farmer asking him to pay 15 lakh, inclusive 7 lakhs incurred for medical treatment of the grandmother. Mr. Y pleaded that he had his parents' jewelry to sell to a maximum value of 4 lakh, which may be adjusted against the dues. Mr. M refused and threatened Y of legal suit to be brought against for recovering the money. Now you are to decide based on the provisions of Indian Contract Act, will Mr. M succeed in filing the suit to recover the money? Elaborate the related provisions. Why? In the case of minor agreements, minor is liable for necessaries. And not only that, quasi contract says the person whoever supplies the necessaries to a minor or an unsound mind or a person dependent on them, for all that I can recover the money. So in this case, can I recover the money? Answer is yes, provided to an extent of the estate I own. So here, what is my property value? My property value is 4 lakhs. Beyond that, minor will not be liable. In this case, whether Mr. M will succeed in the legal suit, answer is no. He's major. For 21 years, sir. All mental health. Sorry. My bad. Okay, my mistake. I repeat wrong. I thought minor. Okay. Mr. M will succeed in filing the suit to recover the money?
Yes or no? Now tell me, good.
Sir, that also no, sir. That time also.
Why?
Like, it's not mentally balanced, no, sir.
Mental
Void contract.
contract is void.
Because with the unsound mind, we can't.
Initially only unsound. What can you do?
Yeah, it's, you know,
People, unsound mind correct only. Then in quasi contract, what did you say? No. You said unsound mind person, you cannot enter into a contract. No. Quasi contract, then what did you see? That is the first one. Law gives me a right. I know. As per law, I cannot. I cannot get back the money. That's why it came under exception. Agreed? No. That's what. So the case will come under quasi contract only. Claim for necessaries supplied to a person incapable of contracting. So all these people will come here only. Minor will also come there. Unsound mind person also will come there. Not only them, even the dependents upon them also will come there only. Yes, sir.
how much you get, sir?
That's what. Read. What does it say? Mr. M supplied the food and other necessaries to Mr. Y, who lost Mr. Y's grandmother. Hence, Mr. M will succeed in filing the suit to recover the money. Now, what is this? Because he's not a minor.
Sir, but he's
The capacity of necessities, that is wherever the estate comes into picture, that will always be restricted to the minor's case. Now, whenever this person has an opportunity to earn it back, minor can be not ratified. We did not say that's for a normal person, right? Can you become a sound mind in the future? Oh, yeah? I'm saying minor case is a dead end. Unsound mind case is the open case.
the not if that something.
Something. that I don't know. something means what? Okay. Okay, let us imagine if this person was a minor, then how will your question change? If it's a minor, I can still recover necessaries, yes, but not beyond estate. Even for necessaries, I cannot recover more than 4 lakhs. Okay. What is the maximum amount of money that can be recovered? Shall the provision of the above apply to the medical treatment given to the grandmother? Hello? So we saw even the person dependent upon them. For them also I can recover it. Answer is yes, no. I can recover. In fact, you remember when we are doing this case only I told you. We can recover. Agreed, huh?
So like you can claim the full amount.
Where?
Okay, up to 3 lakhs you can claim.
Supplier. No, see in this case what they have given. How much is the money he has? The gold, how much he has? 4 lakhs. Now, if you read the question, they have one more information also. What else they have given? Y and his grandmother live in the house. One second. Where is it? Yeah, they live in the house built by his parents. Then whose property is that? Now, isn't it an asset? Can I recover? Yes, I can recover. Why can't I recover? See, what they have, I can recover. I have, okay, see, I have gold. I have property. Gold value they have given you 4 lakh. The total money I need to pay what 15 lakh? Huh? No, 15 includes 7 lakh.
Sorry, plus 15.
Hey,
Total 15.
inclusive. Correct? Huh? Now what they have given 4 lakh gold. Can I sell it and get the money? Answer is yes. I can sell and get the money. Now can I sue Mr. Y for more than gold? Answer is yes. Why? I have property. Yes, sir. Hello. Because in the question they have given the provision. I have the property. Okay. I mean, let us avoid confusion. What is the confusion? First question is, okay, let us take it this way. Minor also leave it. Let us take quasi-contract case only. Whenever you are a person who is incapable of entering into a contract, you're incapable.
Now this person can be minor, unsound mind, whatever. Check the question whether has there been any property given. If property is there, to the extent of property, you are liable. If property is not there, then you are not liable. In my case, I had property. Don't only look at gold. Even house is also a property. So will M succeed? Answer is yes, because money is there, property is there. Sir, let us imagine only gold was there. There was no property. How much can I recover? To the extent of the gold, I can recover. Beyond that is a loss. Again, I repeat, to the extent of gold, I can recover. Beyond that is a loss. In the given case, you have to give given. Now, for example, you can also ask a question. Sir, we do not know the value of property. Yes, write an assumption. Assuming that the property can be adjusted towards whatever is the outstanding amount. Yes, Mr. M can recover the money from 5. Assumption, because they have not given me the value. What else you want me to do? I have to write an assumption. Now in exam, at times, such scenarios may come. You will have to write an assumption. If you look at also somewhere, they would have written an assumption. And rest from the house of Y's parents. See, assumption. Y has inherited the house property on the death of his parents. That's an assumption. Why? Now you look at it. Why they are writing it that way? They're telling Y is living in that house. What if the parents have sold it to someone? That can also happen. That's why they are writing it with an assumption. You also write it. It's valid. Agreed? Tricky itto adike. Understood? Hello? Clear? Same thing is coming. Oh, same. Ricky is the owner of electronic shop. Prisha reads the shop to purchase an air conditioner whose compressor should be of copper. As Prisha wanted to purchase the air conditioner on credit, Ricky demanded a guarantor for such a transaction. Mr. Shiv, a friend of Prisha, came forward and gave guarantee for the payment of air conditioner. Ricky sold the air conditioner of a particular brand, misrepresenting that it is made of copper when it is made of aluminium. Neither Prisha nor Mr. Shiv had the knowledge of the fact that it is made of aluminium. On being aware of the fact, Prisha denied payment of the price. Ricky filed a suit against Mr. Shiv. Explain with reference to Indian Contract Act whether Mr. Shiv is liable to pay the price for the air conditioner. Why? Provision. Sale by description. Correct? Yes or no? Hello? Correctly write down. 1 second. Ricky is the owner. Prisha is the buyer. Shiv is what? Surety. What is the question from? And they're telling you Indian Contract Act. Macha, it is a deception. However you guys answered, everyone answered the same in the exam. Sale by description. No, I'm telling you, that's what people wrote. That's why tricky. Understood? Hello? Everyone fell for it, including us. Yes? What is the question? Question is people. When will agency, when will surety's liability come to an end? Yesterday I told you, reference case. I told you one person, senior asked, go get some reference. Why? Because he had done some embezzlement, I told you. Bills and all he had changed. So people, if creditor conceals or misrepresents any fact, then the surety's liability will come to an end. On those grounds, I'm telling you, whether Mr. Shiv is liable, answer is no, Shiv is not liable. Because not of sale of goods act, it is because of surety. That is nothing but people misrepresentation or concealment of a fact. So surety is not liable. Shiv is discharged from his liability. That should be your answer. No, but that's why understand why I'm telling you see more questions. The way you look at it is changing. That can happen only with questions. That's the beauty of questions. Okay. A bails his jewelry with B on the condition to safeguard it in a bank safe locker. However, B kept it in a safe locker at his residence where usually he keeps his jewelry also. After a month, all the jewelry was lost in a religious riot. A filed a suit against B for recovery, referring to provisions of Indian Contract Act state whether A will succeed. A will succeed by read completely an answer. Correct. He kept the jewelry wherever he would keep his jewelry. He has taken ordinary care. However, I would treat my goods. I've treated your goods also in the same way. And if I still loses it, am I liable? Liable or not? Hello? Exactly. Whenever there is an instruction, it is your duty to follow the instruction. What is the instruction here? Macha, instruction is when there is an instruction, you do not follow an instruction, any liability, you will be liable, even though you have taken sufficient care of the product, even though you have treated the product as if it's your own. Wherever you have kept yours, you have kept that person's gold also there. I do not deny, but there's a specific instruction. If you do not follow, the risk is on you. Understood? Huh? Yes, sir. Exactly. Whatever you said, same only. For a reason they have said that is a bait. They want you to fall there. It's a trap. Wherever I kept mine, that is where it is kept yours also. It's a trap. Understood? Huh? Miss, what is it? Miss A delivered her old silver jewelry to Mr. Y, a goldsmith, for the purpose of making a new silver bowl out of it. Every opening, she used to receive the unfinished goods, silver bowl, to put them into the box kept at Mr. Y's shop. She kept the key to that box with her. One night, the silver bowl was stolen from that box. Was there a contract of bailment? Whether the possession of the goods, actual or constructive, delivered, constitutes a contract of bailment or not? Huh? Bailment, not a bailment. Not a bailment, why? The key was with her. The answer you guys will write it as, remember, the custody was alone given, not the possession. Because the control of the silver bowl is still with her. The key is with her. The bank locker, I told you. So based on that, even though the possession is with him, the custody alone is given with that particular shopkeeper. The control is with me. I am deciding when to open, when to close. That's why custody is given, not the possession. On that grounds, can I claim liability? Answer is no, I cannot claim liability. Why? It is not a contract of bailment. Because control is still with me. Hello? Mr. Ahuja of Delhi engaged Mr. Singh as his agent to buy a house in the West Extension area. Mr. Singh bought a house for 20 lakhs in the name of a nominee and then purchased it himself for 24 lakhs. He then sold the same house to Mr. Ahuja for 26 lakhs. Mr. Ahuja later comes to know the mischief of Mr. Singh and tries to recover the excess amount paid to Mr. Singh. Is he entitled to recover any amount from Mr. Singh? If so, how much money can be recovered? Can anyone share this question PDF? Madhu, I'll share you. I'm adding after the last day, I'll share you. Understood? Question answer, sir. Ahuja of Delhi engaged Mr. Singh as his agent. Ahuja has appointed Singh as his agent to buy a house. So he has asked, can you please buy a house for me? Singh said, okay, it seems. Mr. Singh bought a house for 20 lakhs. So first he purchased for 20 lakhs, it seems. How did he purchase? He told his friend, Macha, do one thing. Go there and purchase this home for 20 lakh. Okay.
and then purchased it himself for 24 lakh. From nominee, he transferred it to his name for 24 lakhs. He then sold the same house to Mr. Ahuja. He said, sir, I have one property. If you want, you can buy that. And he sold it for 26 lakhs. They are telling you, Mr. Ahuja later comes to know the mischief of Mr. Singh. Singh did all of this. They're asking you and tries to recover the excess amount paid to Mr. Singh. Is he entitled to recover any amount from Singh? If so, how much? How much can he recover? 4 lakh, 2 lakh, 6 lakh, or he cannot recover at all? Wait a Pramod.
Like he's property is in name of the master.
The property is in the name of Singh, and that's what he sold. So can he recover? No. What did I do? I did not do any fraud. No. First thing, the agent cannot make secret profits. You are supposed to disclose and make. Why did you do all those transactions? Why? Why? Conflict of interest. Doing interest against obligation. You're buying me a house, but whatever is giving you profit, you're making that and giving it to me. So what is the profit he made? The first house was purchased for 20. You sold it to me for 26. 6 lakhs. I can recover from the agent because it's a, what is that? Secret profit. You're not supposed to make it.
But the
Provision. Huh?
property is in name of city.
Correct. Very good. Property is the name of the thing. How did you get it? Isn't that a fraud? Why did you not directly buy it for 20 lakhs and give it to the principal? Why? So you know you are doing fraud, no? Then agreed, huh? See, logical if you try to see it, will not work. Yes? Okay. ABC Limited sells its products through some agents, and it is not the custom in their business to sell the products on credit. Mr. Pinto, one of the agents, sold goods of ABC Limited to Measures Perul Private Limited on credit, which was insolvent at the time of such sale. ABC Limited sued Mr. Pinto for compensation for the loss caused due to the sale of products to Measures Perul Private Limited. Will ABC succeed in its claim? Answer is yes, because you have to always follow the instructions. If instructions are not there, you have to follow the custom. It is clearly given that in that trade, there is a custom of not selling the goods on credit. So if you sell it, you are selling it at your risk. And that too, you have sold it to a person who is insolvent without acting in due care. There was a negligence. On that ground, yes, I can recover the money from the agent. Understood? Yes, provisions. Focus on provision. Yes. Sonal went to a jewelry shop and asked the sales girl to show her diamond bangles with the ruby stones. The jeweler told her that we have lot of designs of diamond bangles, but with red stones. If she chooses for herself any special design of diamond bangle with red stones, they will replace red stones with ruby stones. But for the ruby stones, they will charge an extra cost. Sonal selected a beautiful set of designer bangle and paid for them. She also paid the extra cost for ruby stones. The jeweler requested her to come back a week later for the delivery of those bangles. When she came after a week to take delivery of bangles, she noticed that due to ruby stones, the design of the bangles had been completely disturbed. Now she wants to terminate the contract and thus asked the manager to give her money back. But he denied the same. Answer the following questions as per Sale of Goods Act. State with reasons whether Sonal can recover the amount from the jeweler. What would be your answer if the jeweler says that he can change the design, but he will charge extra cost for the same? First of all, first question, state the reason whether Sonal can recover the amount from the jeweler. Can she recover? On what grounds? Agreement to sell. So remember people, today we have entered into a contract to buy a jewelry set. Today we have entered, but the ownership will be transferred in the future date, like a carpenter making the furniture. When will the ownership transfer? When the product is complete. This is a future goods. So what we have entered into is called agreement to sell.
Agreement to sell. In agreement to sell, ownership does not transfer when you enter into an agreement. It's a future contract. It's a future goods. So when will the ownership pass? Ownership will pass in the future when the products are manufactured, acquired, owned. Remember that future goods. So in this case, I am not the owner yet. The owner was still that particular jewelry shop person. Yes, sir. Now, on the day, if at all the goods are damaged, the risk is with whom? The risk is with the shopkeeper only, the seller only, not the buyer. So that is the reason. It's an agreement to sell. Ownership is with the seller. The risk is on him. The compensation will be on him only, not on the buyer. Second one, what would be your answer? The jewelry says that he can change the design, but he will charge extra cost for it. This is okay. No, people, it is your mistake. I am not the owner yet. The rectification or damages, you can do it, provided the cost cannot be charged extra. Buyer is not liable to pay. It is on the seller only. Hello? Pakka? Correct, huh? Summer was in search of a second-hand car. For this purpose, he approached Carwala 007, a dealer in pre-owned cars. The sales manager of Carwala showed him the 3 cars which were standing in the parking lane just outside the office. Summer finalized red Wagoner car. After completing the documenting formalities and receiving the price of the car, sales manager of Carwala handed over the key to Summer. But when Summer was coming to parking area for picking the car, the electric pole, hours only. Electric pole fell on the car, which badly damaged the car. Summer claimed that repair expense of the car should be borne by Carwala 007 as car was not delivered to him. Referring to the provision of the Sale of Goods Act, state who will be liable to get the car repaired. Sellara buyera. Sellara buyera. Pramod, you tell them. Why da?
The car, goods is not delivered now, sir.
Not yet delivered. Correct, huh? Now wait, wait. Now Pramod said goods is not yet delivered. Now we'll ask one question to Pramod. Pramod, what are the types of delivery?
Like,
Types of delivery. Actual delivery, symbolic delivery, constructed delivery. What do you mean by symbolic delivery, Pramod?
like they're giving the
They giving?
transfer of ownership to the RC. They have changed the RC.
Correct, correct. Now can you say giving the?
Giving the car key or sir, but he'll take the car.
Pramod is so good. He only knows. He's still arguing. Understood? Provision. Symbolic delivery. He cannot say, I've not yet taken the car. Then what? I should take crane and put it on you. Yes, sir. Delivery is complete. Hello. They have written you, right? Symbolic delivery is good enough. They have just written there are different types of delivery. They have not explained. Some good student has written. Okay. Ayaba. Yenna macha idu? It is like a BCom answer. Okay, read. Punishment alva idu. PTC hotels in Bombay decided to sell their furniture by auction sale. Macha. Oh, idrada. Surprise. Macha, shake. And remember, somehow I have a very strong feeling. This can be an exam question. Yes, sir. Not even once it has been asked. PTC hotels in Bombay decided to sell their furniture by auction sale. For this purpose, they appointed RN Associates as an auctioneer. They invited top 10 renowned architects in Bombay for bidding. A right to bid was not notified by them. Furniture was put up in lots for sale. It was decided. No issues. It was decided that for every lot of furniture, there will be a reserve price. On 25th February 2024, the auction sale was started at 10 a.m. in the lawn of PTC Hotels, Bombay. For a special lot of furniture, 3 parties came for bidding. Mr. Neil Raj Dev on behalf of their respective companies. Bidding was as follows. Neil 5.7, Raj 4.85, Dev 6.10. The sale was completed in favor of Mr. Neil by R.N. and Associates by fall of hammer. Mr. Dev's bid was rejected on the grounds that the right to bid was reserved and the company of Mr. Dev was not invited to bid. For another bid of Italian furniture was made by two parties as follows. Mr. Deer 15 lakh, Mr. Madhu 15.2 lakh on behalf of RN and Associates. Sale was completed in favor of Mr. Deer instead of Mr. Madhu. Mr. Dev and Mr. Madhu argued that the auction sale was not lawful. Give your opinion with reference to provision of Sale of Goods Act. Whether the sale will be considered lawful or not. It is not lawful. Understood the question? It has literally crazy every facts. Auction sale, not even once they have touched these topics. Not even once. Yeah, I'm telling you the history for I can say 10 years. Not even once these points are touched. So remember, somewhere in the near future, this can be a question. Yes. Okay. See what it is. What are they saying? Something and all they said, no? Recomplicatedly written, right? Yeah. Okay. Let us try to dissect. What are they telling? They have written here with a few assumptions. The answer, I wouldn't say it is completely perfect. They have written the answer with a few assumptions as well. But let us try to understand what they are trying to say. PTC hotels decided to sell their furniture by auction. Okay, for this purpose, they appointed R&, Associates as their auctioneer. If you see, someone from R&, Associates is participating in the auction, correct? Somewhere else also he came. Okay, somewhere, I forgot. Okay, see, R&, Associates. Favor of Mr. Neil, correct? So it is clear. Just now I explained you also what? In the case of an auction, seller or anyone on their behalf, if you want to participate in the auction, remember you need to reserve the right to bid. Now, the only question you will be answering is if the reservation of right to bid was made, then yes, this is a lawful auction. If there was no reservation of right to bid, then it will not be a lawful auction on that party. Now, what we need to check is, did RN and Associates, did they reserve the right to bid? We need to check whether any information like that is given or have they specifically given that there is no right to bid. Was not notified, then that's all people, whatever RN Associates, in our case, they are given something. Who represented RN Associates? Madhu. So Mr. Madhu argued that auction sale was not lawful. So we will say, no, it is lawful only because the right to bid was not reserved. That's why they rejected your bid. That's what was the problem, right? See, in the second case, what happened? Dheer has given it for 15 lakh. Madhu has given it for 15.2 lakh. Sale was completed in the favor of Mr. Dheer. Madhu is telling whatever you guys did is unlawful. We are saying no, what we did is lawful only. Because you guys did not reserve the right to bid, you cannot participate. That's what I'm taking the stance. So my rejection is lawful. Huh?
If they reserve the right for bid, if it is not lawful.
Yes. That's what I told you in the auction sale. No. An auctioneer, if they want to participate in the bid, imagine, I think it's a very good, valuable furniture. I can sell it for a higher price in the future. I can also participate, disclose and participate. Just like agent, don't make secret profits.
Bid one is for bid it for 50. If they bid it for 20 lakhs, finalize Deal bid it for 20 lakhs.
Deal for 20.
15.2 lakhs.
15.2. You tell me, whenever you're selling a furniture, I'm selling my mobile. Will I sell it for a higher price, lower price?
higher price, no, then I will definitely go with 20. That was the problem with Madhu also. Dheer has given 15. I have given 15.2. They have rejected my sale. They have agreed 15. That's why Madhu is saying whatever you guys are doing, it is unlawful. They are notified. Then I can participate. Then I'm clearly told, no, that even I will be participating like one amongst you. I'm clearly telling it and doing that. Then yes, it is valid. It is given in the law only. Then yes, I can do. No problem. Agreed. All of you. And the next one now. What is the other question they have? Mr. Dev has a problem it seems. Why? Go back and see the other one. They invited the top 10 renowned architects in Bombay for bidding. A right to bid was not notified by them. Furniture was put in lots for sale. It was reserved at every lot of furniture with reserve price. The auction sale was started 10 a.m. in the lot for a special Neil Raj Dev. Dev came on behalf of respected. Bidding was as follows. Mr. The sale was completed in favor of Mr. Neil by RN and Associates. We gave it to him, it seems. Is it valid? Of course, it is invalid. They have represented on behalf of. Correct, huh? Mr. Dev's bid was rejected on the grounds that the right to bid was reserved and the company of Mr. Dev was not invited to the bid. So they are telling you the right to bid was reserved and the company of Mr. Dev was not invited to the bid. What are the grounds they are telling you people? In this particular case, they have taken no, in this case, they are telling you that they have reserved the right to bid. In this case, they have reserved the right to bid. If they are giving you, take they have reserved the right to bid. If they have not given you, don't take that they have a right to bid.
So, if they say buy R and associate, it means that they are telling that they are the auctioneer, so they did the auction. It doesn't mean it's on behalf of them, right? Mr. Neil buy R and associate means the auctioneer has selected Mr. Neil. Because they was not invited.
Have they given that he is representing R and Associates somewhere? They have not given.
Only Madhu is represented, and they.
Mr. Neil, Raj, and Mr. Dev. The sale was completed in favor of Mr. Neil by R and Associates by fall of hammer. Yes, whatever you said is right. They are not telling that Dev is representing on behalf of RN and Associates. They are telling you it is two different sentences.
Sir, but the auction is closed.
That I come back and tell you. So, no, the confusion was, see, she was confused. Why is it considered as valid here? Why is it considered as invalid here? RN and Associates representative only bidded in one place, not in both the places. This part is clear. See, I thought they are representing someone from RN Associates even in the first case. Answer is no. Neil, Raj, Dev, none of them are from RN Associates. In the second part, one person is participating on behalf of RN and Associates. Second case, they are participating on behalf of RN and Associates. Second case. And that is why in the beginning they have given right to bid was not notified. On those grounds, the second sale is whatever they are trying to tell. That is, yes, RN Associates cannot participate because right to bid was not reserved. In the first case, what is happening? There are three people who has participated. Who are they? Neil, Raj, Dev, on behalf of their respective companies. Now they have auctioned accordingly. The sale was completed in favor of Mr. Neil. Who completed this sale? They're telling you it was completed by RN and Associates. That means that's a company who said yes 3 times fall of hammer. They said Neil won the bid. Agreed? Okay. And what they're telling you? Okay.
Let us keep it clear. Okay. Now see what they are telling you. Now see here. The sale was completed in favor of Mr. Neil by RN and Associates by fall of hammer. Mr. Dev's bid was rejected on the ground that the right to bid was reserved and the company of Mr. Dev was not invited to the bid. The company of Mr. Dev was not invited to the bid. Now the question is, people, somewhere in this entire question, has they given anywhere, have they mentioned in the question that it is an open auction or closed auction? Have they given? I'm asking you, you see the question and tell me. Okay, so then I tell you two interpretations. We are conducting an auction. We invited 10 people also to the auction. Specifically, please, you also come. Second interpretation, please only you 10 come. It is not open for everyone. I'll give you two interpretations. One, auction is open. I'm calling you 10 people also, please come and participate. First interpretation. I'm giving invitation, please come. Interpretation number one. Interpretation number two, only you 10 people come for the auction, no one else. We have invited only you 10 people. If you ask me, is that part clear? Answer is no. They have not clearly given. Have they given that? Have they given? No, see, even I am also seeing it now only. When I saw it, I saw the question, I just copy pasted it. That's why even I am seeing. Read it. If you find any word, then it was a closed bid. If it was given somewhere,
Their bid was rejected on the ground that right to bid was resolved. The company of Mr. Dev was not invited to bid.
Mr. Dev was not invited to bid. That's what I'm telling you. We did not invite Dev to bid. Now my question is, was it an open auction, closed auction? Closed auction? Yes. Now people, now that's what I'm saying. Why I'm saying that is, I tell you why. Now come back and see your answer here. In the first auction said the rejection of Mr. Dev bidding was not justified since the information as to right to bid was not expressly given. That means what? They are taking an interpretation that whether it is an open auction or closed auction, that information is not expressly given. They have taken that interpretation. Is it valid? I would say the question is unclear. If you ask me, the same thing comes, write the same thing and come. They have taken it as an open auction. They have assumed it that way. That's why I'm saying, even see what you're feeling is correct. Because it is a playing of letters. We invited only 10 or we invited also 10 people. It's an interpretation problem. We will interpret this way, they interpret it that way. But what you felt isn't correct, answer is 100% yes. See, exactly I'm saying what you feel is correct. I will tell you the other part also. If I was a student, even I also would have written, it is a closed auction. Because I always tell you, there will be hints. That these are hints is what I will say. 100%. Now I'll tell you one more thing also. Not every answer given by the institute is right. Yes, sir. That's why they say these are all suggested answers. So not every answer given by the institute is right. In the past also it has happened. Answer is wrong. Yeah, we can take that. But why am I not telling you here this answer is wrong? Because I gave you that interpretation. You got it? We invited 10 people for the bid. It can be like, it's an open auction. And we are giving 10 people also. We are calling them also. That is also okay. For example,
There is marathon. ICU people are there? People apart from ICU? Anyone from outside? Now see, there was an invite. There are 3 set of audience here. Now this marathon is for whom? Exactly. In the auction, we invited outsiders. You can come and attend. We called our students. We called ICU people. Now who exactly are we calling? Now when I called only ICU, can I say is it only for ICU? Exactly what I'm trying to tell. They're telling we invited 10 people also. We invited ICU also. What you're saying is 100% correct. But take it the other way. What if I feel you will miss out coming to this auction? I want you to be there. Can I invite you? Like a special invitation? Because we know not everyone can buy. Worthy people who really can afford, I might have called them. But that doesn't mean I will close doors for others. That's an interpretation, absolute interpretation. Getting the point? Now, what you felt is 100% correct. Now, when there is a, now your question is, sir, what to do if this question comes in exam? Suggested answer, write it. Cut copy paste and write it. That's why I took it. If this was not taken in exam, we will write the other way around. Now we can claim it because you said it is a suggested answer. If we write the other way, we can't claim it. Agreed? Yes, just like KVA tempter, exceptions to KVA tempter, Sale of Goods Act. I'm telling you, patent or brand name, I'm telling it for the last 7 attempts, it is wrong. But it is still written under exceptions to KVA tempter. Then it is wrong. That's all. Wrong. Hello? Pakkana? Yes, sir.
We just like we're assuming that it's a closed.
Write an assumption. No. If you write closed offer, then the answer will change. Here they are telling you, nowhere it is mentioned that an outsider cannot participate. So the rejection of Dev's bid is invalid.
We can say that Dev's bid was invalid and say that Mr. Neil is valid.
You're saying first case, huh? Neil only won it, no? Huh?
Dev's bid was slightly rejected.
Who won the bid?
Neil got won the bid and the sale to the Neil was accepted.
Valid.
Both the case, sale to both are up.
So second case is unlawful.
Second one is unlawful. Second one, there is no doubt, no?
No, second one is unlawful.
No, I didn't get your question. Second, are you combining first and second?
Saying both are up. Sale also was lawful. In that case, we can reject the Dev.
Dev is rejected. That's what we saw, huh?
The Neil won the bid.
Correct, yes. Highest bid.
It's lawful.
No. See, what they're telling you is, if at all you did not reject Dev's bid, then who would have won? Then how can Neil win? Dev has bidded for 6.1 lakh. Neil is 5.7 lakh. And what Dev is trying to tell is, you have unlawfully rejected my bid. Now they're asking you what Dev is feeling. Is it right or wrong? The answer that is suggested is they are telling you what Dev is feeling. That is right. You have not lawfully rejected. You have rejected it unlawfully. So if you have unlawfully rejected, that means can Dev participate in the bid? Yes. How much is bid price? High or low? Then who should win? Neil. Then will he win? No. Understood? Got your point? But if at all, if Dev's rejection was lawful, then yes, Neil will win the bid. Exactly what happened in the second case, no? RN and Associates have bidded for highest 15.2. We rejected them because right to bid was not notified. The next highest bid was 15 lakh. That's why you won. That was lawful. That's fine.
but the first one was not lawful. They've had a right to participate in the bid, but you wrongfully rejected him, is what they are telling you. Hence, it is unlawful. Second one is lawful, first one is unlawful. Correct, huh? They should not have rejected. First one they have rejected, it's good. Clear, huh? Hello? A very different perception. Trust me, till today auction, they have not done this. Yes? Okay, good. Something I hope you guys understood. Okay. Okay. We'll go back, huh? Online, whatever you are saying is 100%. Hey, I am not the advocate of ICA's answer. I'm telling what else you want me to tell. That is a suggested answer. I see. I can tell you people it is wrong. Write whatever I'm telling. If you lose a mark, you will come and question me versus you questioning ICA. Which one will be valid? You are. Hey, where will you and me go? Better to question them because you're writing on their answer. Again, I'm telling you, what you said is correct. Even if I was a student, I would have written the same. It's a close bit because so many places there are hints. Even I don't know. See, I cannot call it out because it's a recent one that I've taken the question from. Until you have a conclusive thing, I can say it's a mistake. It's wrong. It's 100% wrong. Yeah, but they have suggested it as an answer. And why I'm telling that is at least in one place that there can be an assumption that it was an open auction or it's a closed auction. It's an assumption that they are writing. Clear, huh? Hello?
If the right to bid is reserved, that one we can consider in case of anybody, like auctioneer, seller. Not both the cases because in textbook it's only for seller. Right?
Seller or any other person acting on their behalf.
But that one.
So, for example, BCCI wants to sell people, auction people. BCCI won't sell, no? They will appoint that middleman. Now, that person will come and sell. Now, they are not our, what is that? I mean, they are not, Ganguly won't come or JK Shah won't come or, sorry, JK. Sorry. Yaar guru number? Amit Shah, sorry. Jay Shah, sorry. Okay. Yes, sir. So, so I cannot say that they are appointing someone else as a middleman.
Example of that clock example.
Ah.
Those people really like it because they only wanted it. What RNS associated really like the furniture, they only wanted it, so they put for it. And if the right of bid was reserved for the seller, it means the main company, anyone on behalf of them cannot bid. But Madhu can bid on behalf of RNS associates. If the right to bid was reserved only for seller.
No. So you can take it in both the ways. It can be reserved by the seller directly also, or any person acting on his behalf. Let it be even an agent.
But Madhu is not acting on his behalf.
On whose behalf? RNS associates, sellers associates. On sellers' behalf, they are not acting.
They are RNS associates.
Correct.
They like the furniture. They want it for RNS associates.
You're saying an indirect way. I didn't get you.
So the clock example you gave. They like the clock they wanted, so they wanted to bid.
RNS associates, you're saying.
Sir,
The auctioneers, you're saying. Auctioneers wanted the clock.
they wanted to bid. So
Hmm.
if the right to bid was not reserved, they could bid.
Who could bid?
Auctioneer.
No. They can only bid if they reserve the right to bid. Because now imagine, I am a neutral party. If I am only coming and participating, that means it will be unfair. I would have had some advantage. So if even the seller, it can be auctioneer, even if he wants to come and participate, it is his duty to come and disclose that I have to reserve the bid.
Only then even the auctioneer can also participate.
Very important. It's our other person actually.
Seller is other person, auctioneer means? Auctioneer has to act on behalf of seller only, no?
The option also there is.
No, see. In auction sale of lot 2, since right to bid was not notified, it shall not be lawful for the seller to bid himself, to employ. So it can be the company itself. Now, who is coming on behalf of the seller? Auctioneer. Now, they can also not bid until they do not reserve the right to bid. So, on this case, yes, the rejection was lawful. Yes. Clear? Huh? Hello. Okay. Chapter 1, Taka we do out of Indian Partnership Act 1932. General nature of partnership da. Definition of partner. What is partnership da? Relationship between persons who have agreed to share profits of business carried on by all or any of them acting for all. So any of them acting for all or all of them acting for all. This concept is called as what? Mutual agency. So if one partner goes and signs the contract, he is binding all the other partners in the partnership firm. Agreed? Huh? Yes, sir. This concept only is called as mutual agency. Elements of partnership, there will be 2 or more person. That can be artificial person or it can be natural person. But remember, a minor can be a partner. Huh? Minor cannot be a partner. Minor can be a beneficiary. What is the maximum number of partners in partnership? 50. The maximum number of partners in partnership firm is 50. Where is it written? It is not. It is written in.
Association for any association.
It is written in Companies Act. According to Companies Act, any association of person which is going as unregulated entity, you cannot have more than 50 people. If you go beyond 50 people, it will be considered as illegal association according to Companies Act. So according to that, the maximum number of partners that can be there in partnership is people. Next one, business. There has to be existence of a business. Meaning what? There can be a question here. You cannot run a non-profit organization in the form of partnership. Like we have Reliance Foundation, Infosys Foundation, Isha Foundation, all these foundations are there. They cannot exist as a partnership. They can exist as a company, trust, society, but not as a partnership. Why? Partnership in India has to earn business. That's the definition, no? Yes or no? Who have agreed to share profits of business. Business is clear, no? It cannot be not for profit. No. Hello. Cut, copy, paste applies to LLP also. You cannot run a LLP for NPO activities. It should be for profit. Hello. Somewhere important. They can ask you in the form of partnership or LLP. Answer is same. You cannot. It has to be for business only. Next one. Agreement to share profits. Can one partner take all the profits? Can one partner take all the losses? Definition says it's a agreement to share profits. Definition does not have losses in it. So a partnership, one partner cannot be entitled for 100% of profits. A partnership cannot exist. But one partner can take 100% of losses because definition does not stop it. Remember and go. Hello. Business carried on by all or any of them acting for all. Nothing but mutual agency. True test of partnership agreement. Meaning partnership is created by agreement and not by status. What is this? Not by status. HUF. By birth you become a member. No. But here you have to become a member by agreement only. Sharing of profits of business. Remember, in many cases you will share money, but not every sharing of money can be considered as sharing of profits. For example, employer will pay money to employee. Can I say sharing of profits? It is a remuneration. Correct? No. You pay money to your bank for the loan you have taken. Can I say that? Imagine I started a business. I took money from a bank. Can I say he is my sleeping partner? Any loss happens, catch the bank also. Can I say, see, I'm praying every month, I'm paying him money also. So what am I paying him every month? That is considered as interest and not considered as profits. So there will be sharing of money in many cases, but not everything can be considered as sharing of profits. A partnership firm, imagine there were 3 partners. One partner dies. Out of goodwill, the other 2 partners agreed to give a monthly maintenance to his family. The family is claiming that we are partners in the business because we are getting monthly pension. Can I consider it as sharing profits? No. That's what I'm saying. There will be sharing of profits in sharing of money in different names, but not everything can be considered as sharing of profits. Remember, they will give you this exam. They will ask you. They will give you 4 or 5 scenarios, and they will ask you, does this amount to partnership? These are the examples. It can be receipt of money by lender, that is bank. What the money we give them, it will be called as interest. It is not sharing of profits. We giving money to employee, servant, agent, you will treat it as remuneration and not as profit. Same thing, receipt of annuity, pension to a widow or a child. It is a monthly maintenance. It's a pension. It is not sharing of profits. Hello? Most popular one is this. Some 8 times they would have asked them. What do you make co-ownership of? A had one property. A has 2 children. BA, CA. A died. The property, there are flats in the property. Rent is coming. The rent is equally split between B and C. Now the question is there any partnership between B and C? So remember, it's not a business. You're not using your brain to do something there. Automatically money is coming. You're not using that particular thing as a business. There are no decisions made. There is no business that has taken place. Then what do we call such things as? We call it as co-ownership. It's just the rent that you're getting. You cannot call it as partnership. Hello? Pakana. And the last one, receipt by previous owner as a consideration for goodwill. What do you mean by that? A person who has left the business, we have paid him some money as a settlement. We have given that money. In some cases, they will still give for 1 year, 2 years. They will give money. They will keep on giving money. For example, I forgot the movie name. Netflix was giving a share of profits for the movie being sold on Netflix. Because of that movie, whatever revenue Netflix was making, it was from some Hollywood movie. Yeah, they filed a case when this particular agreement was stopped. Now imagine my movie is listed on Netflix. Netflix is giving me money for say 1 year. Can we say that there is partnership between us and Netflix? No. For selling the product as a matter of goodwill, they have agreed to share some revenue for a certain period of time. I cannot consider it as profit. I cannot consider it as partnership. That is only called as goodwill. Hello? You getting it? Okay. Next one, mutual agency. True test of partnership, section 6. That is, if at all there is, what is that? A partnership should exist. These are the 3 things that you guys need to check. Only these 3 are, sir. It depends upon case to case. A court, if at all they want to prove whether there is partnership between them or not, they can check more also. They will check whether accounts are there. Have they been registered? Have they maintained separate books of accounts? They can check everything and they can say whether between them there is partnership or not. Agreed? Huh? That is what was given in this case law. Santiranjan Das Gupta versus Dasiran Mursamul. Same thing. The court tried to identify certain aspects and they said whether there is partnership between them or not. Like they said there was no records of terms and conditions, meaning no agreements. There were no accounts maintained, no bank accounts. They were not registered also. Keeping all this in mind, they said this cannot be treated as partnership because there is no evidence of existence at all. Understood? Huh? Hello? Kinds of partnership.
Partnership for fixed period. What do you mean by that? In partnership, we clearly write it will be valid for 5 years. Such type of partnership is called as partnership for. Can I continue after 5 years? In the deed, we have written it will be valid for 5 years. Now 5 years is completed. Can I continue after that? If at all the partnership was for a fixed period, if you continue the partnership beyond that, remember it becomes partnership at will. You can still continue. There is no hard and fast rule that after 5 years you guys have to dissolve your partnership. You can still continue. The partnership will become partnership at will. What do you mean by partnership at will? Will means people, your choice. You will exist until you guys want. If any one partner gives us notice and says, let us wind up, you will wind up. So what is a partnership at will? At will is nothing but at the option of the partners. If they feel it is time, you give a notice that let us dilute, you will liquidate. That is only called as what? Partnership at will. You are existing because of your choice. If you want to wind up, you will wind up. Next one is called a general partnership. What do you mean by general partnership? A partnership which can do under the same name 3 to 5 businesses is called as a general partnership. ITC sells pufu pufu. They sell Sunfeast, no? FMCG products, no? Classmate, no? Everything, no? Yes or no? General partnership. They are not partnership, they are company only. I'm saying you example. If there is one particular thing, they are doing 3 to 4 things under that. You call it as what people general partnership. What do you mean by particular partnership? They are doing a specific business. It's called as. If the particular thing is completed, for example, we are doing a partnership with, say, for example, government for metro. Metro is completed. The project will come to an end. Now it's a private government partnership. After the metro is completed, the partnership will come to an end at their choice. Or no, we want to continue this. Okay, continue. So that's such type of thing is called as what people? Particular partnership. Types of partners, active partner. Who is active? Me. Who is sleeping partner? You. Active partner is a person who actively participates in the business decisions of a company. Remember, whenever an active partner retires, resigns, it is his duty to give a public notice. Your liability will continue until you give public notice. Exam question they can ask you. Sleeping partner, who is he? Sleeping partner, a person who has just contributed capital, no efforts. The world does not even know that this person exists. If he retires, should he give a public notice? Not needed. No one knows. But his liability will always be there. Next one is nominal partner. Who is nominal partner? A person who just gives his name is called as nominal partner. These people are like those who are having some value in the society. If their name is added, then there will be reputation that will be added. They won't do it for money. They do it for relationship generally. But I'm not telling. If you see your books, they say that they don't expect even profits. But that is not the case. You can pay money even to nominal partner also. There is nowhere it is written that nominal partner will not be entitled for profits. If we see our book, they have written it that way. But it is not the case. Nominal partners are also entitled for profits. If nothing is there, then why will they do? Yeah. So nothing like that. They can also be entitled. They are generally what? Celebrities, industrialists, big people. If their names are associated, it is good. That's why we take them. Next one, partners in profits only. Who are partners in profits? Example is minor, but anybody can be partner in profits because one person can take all the losses. That means all the other partners are partner in profits only, no? If there are 4 partners, one partner is taking 100% losses. That means the other 3 partners are partner in profits only, no? Incoming partner, Anana. Outgoing partner, Anana. Partner by holding out, estoppel. Our Nitish case,
Correct? Huh? Partner by holding out is nothing but a person who goes to the world and says, I'm a partner, in front of partners only, and they keep quiet. So you are giving the unnecessary assumption in the mind of the world. Oh, this person is actually a partner. So the other partners should have stopped him. Correct? Huh? Exam question now. A, B are the partners. C is a manager in their firm. Hello? Now, one day B was going to one bank. B asked C, will you also come? B took C along with him to the bank. In the bank, B introduced C as their partner. C did not deny it. C also said, yes, I'm a partner. C also felt happy. So C was introduced to the bank as a partner. So people in the eyes of this bank, C becomes a partner by holding out. This only is called as partner by estoppel. Remember, C is for, let us imagine if A and B does not pay the loan back. If any notice is sent, C will also be liable to this loan. Let us imagine because of this contract, if the partnership firm earns any profit, C is also entitled for that as well. Loss also entitled, profit also entitled. Now, sir, this bank, let us imagine ICICI Bank. The partnership firm did not pay the money, whatever loan they had taken, they did not repay. So, ICICI Bank sent a notice to A, B, and C to repay the loan. Is C liable to pay? C liable to pay or not?
Yes, sir.
Partnership firm has taken loan. They have not repaid. The same ICICI Bank, wherever he was introduced as a partner. Now, because the loan was not repaid, ICICI Bank has sent a notice to A, B, and C to repay the loan. Is C liable to pay or not? Yes, under the grounds of estoppel or holding out. So C recovered. ICICI Bank recovered money from C. On the parallel universe, there was one more bank, Axis Bank, from whom A and B long back had taken loan. ICICI Bank said, A, we have recovered the money from A, B, and C. You also file a notice on C. You will be able to recover money. So Axis Bank also sent a notice to A, B, and C. Is C liable to Axis Bank or not? You got the question? He's a partner, Noda. Estoppel, holding out. Can Axis Bank recover the money or not? Understood the question or illa? Question understood. Can Axis Bank recover the money or not? Holding out, partner. Remember people, exam question now. ICICI Bank, till there we are clear. We are not clear for Axis Bank. Axis Bank cannot recover the money. If at all, C has gone and represented as a partner even in front of Axis Bank, then you can recover.
So new partner cannot be liable for
That I'll tell. No, what he's saying is different thing. I'll tell that. We'll come back that. I'll not take it here. What he said is correct only. But I'm saying I'll not clump it. Now what I'm saying, let us imagine same time the loan was taken. ICICI Bank alone, I was introduced as a partner, not Axis Bank. A person who is not aware cannot recover the money from the partner who is holding out. Wherever I was represented as a partner, only from there I can recover, not from every place. I think Axis Bank cannot recover the money. Understood? Hello? Done. The second unit, sir, relation of partners. Sir. What are the relation of partners done? You have a question, done?
you will probably know that.
Yeah, I will tell you. When we come across assignment, I'll tell you. Transferring. General duties. What are the general duties of partners done? Just to be just and faithful, give true accounts. Duty to indemnify means what? If at all because of you, if the partnership firm suffers any loss, it is your duty as a partner to pay for the loss. Rights and duties of a partner, it is always decided by the contractor. What is your right? What is your duty? It is all given in partnership deed. Correct? Can we revise the partnership deed? Is it possible? Yes, provided all the partners have to agree. You can change it. Agreement in restraint of trade is valid as long as it is reasonable. Meaning what? As long as you're a partner, you're not supposed to be a partner or you're not supposed to work in any other place. Is this restriction valid? Answer is yes, reasonable, valid. Conduct of business. Partner will have to do it diligently. Okay, any differences of opinion? Meaning, whenever we want to decide something, we always decide based upon majority, usual matters. But if at all something very important, like change in nature of business, till today we were doing education. Now let us do, say, finance business. We want to change the nature of business only. If this decision we want to discuss, majority approval will not work, you need to take unanimous approval, meaning all the partners have to agree. Every partner can inspect and take copies of books of accounts. Your thing, except transferee, it will come again. We'll see when we are doing transferees rights. Important. Mutual rights and liabilities. Right to remuneration. Does the partners have right to remuneration? Yes, sir. By default, you are not entitled for remuneration. You can pay. If at all your agreement provides so, you can pay. Even if your agreement is silent. If it is customs. Customs means what? Traditionally, for the last 10 years, we have been paying remuneration. It becomes customary and hence you can pay remuneration. Exam question they can ask you. Yes? Next one, right to share profits. How will you share profits? As per the ratio given in the agreement. If ratio is not given, then equally. Remember, few people will think it is a capital contribution. No, you will always meaning divide it equally if nothing is agreed. Interest on capital, can I pay? You can pay in your partnership deed. If it is written, you are entitled for interest on capital. You can pay. What if my partnership deed is silent? If your trade or customs provide, I can pay. What if that is also silent? If any other statutory provision, if some other act says you can pay, you can pay. For example, Income Tax Act allows you to pay up to 6%. If it is given in some other act, it is given, yes, it is given. So can I pay? Yes, I can pay. Remember and go. Clear? Interest on advances, we can pay up to 6% per annum. Right? I have a right to be indemnified. What do I mean by that? Because of someone's mistake, we all had to suffer the loss. For an outsider, we all will be liable. But amongst us, it is whichever partner did the mistake, it is his duty to indemnify the people who suffered the loss. Understood? Meaning, if any partner did a mistake because of his wrongful act, if we suffered loss, the partnership firm is liable. We have to pay. So, for example, if you ask me, there are 3 partners. A takes care of sales, B takes care of finance, C takes care of operations. What do you mean operations? Manufacturing, all of that. In the factory, all the responsibilities of C. Now, what happened one day? There were big plant and machineries, but they were not properly covered, meaning not properly fenced. Whose responsibility was it? It was a responsibility of C to take care of all of that. But C did not take care of that particular aspect. One of the employee, while working, he was putting something. His hand also went inside the plant and machinery. Yeah. Strawberry juice came. Now, people, you tell me, whose liability it is? A and B are telling, we are not liable. I have taken care of my sales department. I have taken care of my finance department. The employee has filed a case on you. You are liable. It comes under compensation, permanent disability. You will have to pay compensation to the family. Now, who will be liable here? Partnership firm as a whole is liable. But tell me, now who did this mistake? Now that is what they're telling you. Because of you, if any loss happens, let us imagine, I'm just giving you one of a scenario. For the outsider, the partnership firm is liable. But amongst the partners, It is C's mistake. C is liable to indemnify the loss. You have to give the money to A and B. If they suffer anything from their pocket. Hello? Let us imagine A, B, and C. They go and they borrow money from ICICI Bank. C goes and borrows money from ICICI Bank. C takes that money. C runs away. ICICI Bank wants to recover that money from A to B. Can he recover? Yes, yes, you're liable. But Macha, it was your fault. It is C's responsibility to indemnify A and B. That's your duty to indemnify. Agreed? Huh? Okay, partnership property. What and all partnership property can be? Partnership property can commence, meaning partnership property can include what and all. What and all you started with. So at the time of commencement, what and all you brought in, it can be capital, it can be furniture, it can be car. Everything will be considered as partnership's property. What else will be considered as partnership's property? Whatever you have earned during the course of business, meaning after started for the next 5 years, we have added some assets. We have added some land. We have acquired some plant and machinery. That will also become the assets of partnership firm. That's partnership's property. What else is considered as partnership's property? Goodwill. Even that also has some value, right? I can sell it, I can realize it. Agreed or not? Yes, sir. Okay, next one. Personal profits earned by partner. Can a partner earn personal profits? Huh? If you earn, what will happen? You have to say, people, if you ask me, agent, whatever you saw, secret profits you cannot make. That's all. A partner cannot make secret profits. First one. A partner cannot make competing business. What do I mean by that? Imagine if we are into education business, one more partner also cannot run an educational business. Whatever profits he is making there, he has to give it back to the partnership firm. He is liable to give it back to the partnership firm. Any secret profit made or any competing profit made, you have to give it back to the partnership firm. What do you mean by secret profit? Imagine this institute is closed in the night. So one partner comes and runs night classes here. Whether other partners are aware, no. He's running his personal classes using the firm's property. It's a secret profit. One partner goes to an outside world, he will introduce himself. I'm coming from so and so partnership firm. I'm using that name to get some work done. I'm using that influence and I make some money there. It is my duty to repay back to the partnership firm. That's the meaning of if you earn money, or imagine we want some raw materials. I will give the contract to someone. I will charge some commission, 5%. All of this, I have to give it back to the partnership firm. I cannot make these profits. Simple, huh? Next one, liability to third parties. All the partners are jointly liable. We know that. Yes or no? Liability of the firm for wrongful or negligent acts of the partner. What is this? Strawberry juice. Is the firm liable? Sir is yes. Liability of the firm. Who is liable? He acted in his ordinary course within the partner's authority. Agreed, huh? Hello? Liability of a firm for misappropriation. What is misappropriation? ICICI Bank gave loan. C took it, ran away. Is the firm liable? One partner took the money, ran away. Is the firm liable to repay that loan? Yes or no? Da? Pagga. It is firm's liability. If the loan was taken in the name of the firm is liable. It is a duty of this person to indemnify. But is the firm liable? Answer is yes. The firm is liable. Relation of partners to third parties. Partner is an agent of the firm. Implied authority of the partner. What do you mean by implied authority? Da? Authority to bind the firm. For example, I just said C should take care of operations, that is factory. I did not clearly tell C's responsibility is to put fence near the plant and machinery. I did not tell it anywhere. If I tell you need to take care of operations, it is your duty to do everything under that. Agreed? Huh? That is the meaning of implied authority. I'll give you one power. Because of that, you will have to do everything else. Now, for example, to tell you that, now imagine, we will ask Pramod. Pramod, you will have to arrange, say for example, one award function for Arivu. Now you all will pass, no? Say yes, da. Now you all will pass, no? Now for that, you have to organize one award function. What and all you will do. I'm giving you a right and I'm going. Whatever you do, I will take care of it. But you have to organize a really good event. Now tell me what and all you will do. Okay, you'll get a stage, awards, decoration, okay. Food also needed. Food, juice, refreshments, entry drink, exit drink, DJ, create. Gift, gift, cash prize, Papa, day. Green. Voucher. Bouncer. What are you guys organizing? Okay, bouncers. DJ and lights on the auditorium. Honorarium, the play money. Okay, guests and all, okay, guests. That and all, no. Who wants guests and you keep it on table, we'll take it. Correct. And commentators, okay. And singers, okay. Dancers. Acri, ಏನೇನ್ ಆಗ್ತಿರೋ acri and DJ on they said and finally someone says faculty. And a bouquet. Saka. Now I just told him arrange one award function. He did one marriage only. Now my question is, am I liable to pay for all of this or not? I'm liable to pay. If you say so required, sir, are you DJ correct? The people what is it is called as I just told him one word award. I don't know 20 ticks will come with that stuff. But okay, let us imagine if at all to arrange an award function, if you really think all of this is required, now what Pramod had is called as implied authority. I am liable. I did not give him power to do each and every one of it. I did not give him that right. But he did literally everything. Agreed? In every place he will go and say, ArivuPro will come and pay. ArivuPro will come and pay. And he also went and he has also got one new blazer. He has to look good, no? Now he has come and said, ArivuPro will come and pay. Now my question is, you tell me, should we pay? Why? Implied power? Understood? In implied power, you can't bring your friend house and get married. Sir, anyways, all of this is happening. Silent Papa, he'll get married. Implied power has some restrictions. Within the power, whatever we do, the partnership firm is liable. But if you are going beyond the power, the partnership firm will not be liable. Agreed? But let us imagine, now this Papa, that person who gave him blazer, believing ArivuPro will come and pay because we paid for all of these people. What about that person? The law will ask one question. What? The third party is liable or implied authority is restricted when? Now, only question. Does the third party know about the restriction? What do I mean by that? Does the third party know that he can only do these things but not getting a suit? Does the third party know? If the answer is no, then we will ask the second question. The third party does not know that he is dealing with the partner of the firm. Now, the second question I'm asking, does the third party know that he is a partner in a firm or he does not know? They are thinking is Pramod. Pramod can act in two capacities, right? Now, for example, imagine if at all, if Pramod wants to open a, he wants to buy a car, he can buy for him. He can also sign as Mr. Pramod, partner in ABP and Co. Both the places his signature only. But in one place he is buying it for him. In one place he is buying it for the firm. So now we will ask the third party. Did you know that Pramod was a partner in the partnership firm? Did you know that? If they say no, or if the answer is no for both people, then what we will do? We will say that we will not be liable. You please take the cost of the suit from Pramod only, because you neither knew that he was a partner and you also knew that there was a restriction that suit price we will not pay. If you know everything and if you are still giving, you are giving it at your risk. Are you getting the point? Hello? Uh,
That he can't able to buy the suit. Yeah, then who is it?
no, if third party is aware of the restriction, now third party knows that you are not supposed to get a suit. I know that you are a partner, but I know that you cannot get a suit. In that case, the partnership firm will not be liable because you are aware of the fact. If the third party does not know, you are not even a partner.
So no, they know about he is a partner.
Huh. Partnership firm will be liable. Because if the third party does not know about the restriction, then the partnership firm will be bound to repay the loss. Now, we will recover the money from Pramod. Duty to indemnity. Clear? Huh? Hello. Next one, transfer is rights. Much important. Exam point of view. Hey, A, B, C, da. C can sell his share to D. Possible? Huh? Can you sell your share to an outsider? Possible?
Yes, generally no.
So generally no, but I want money. Where do I go? I will first ask A. Hey, will you buy my share? I need money. A says no, no money. I go to B. Hey, I want money. Can you please buy? B says no, I don't have money. Then C cannot be stopped. C can sell his share to D. You cannot stop him because then how will he get his money? Correct? Yes, sir. But remember, when the new partner is coming in, that is Mr. D, he has certain rights, he has certain liabilities, meaning restrictions. What is the right? If D is coming in today, he cannot get the same right as C has, meaning he cannot involve in the decisions of the partnership firm. He cannot involve in management of the partnership firm. What else he cannot do? He cannot get the books of accounts. Then what is he entitled to? He will get the share of profit. That's the only thing he will get. Nothing else he will get. On the day of the winding of dissolution, that day he will get the accounts as well as you will also get the total share of whatever is the part you have. Of that, your share you will get. That is what is the transfer is rights and restrictions. Remember, exam point of view, they can ask a question. Clear? Okay. Next one, the new partner. Kind of, see, that's what interfere, require, only entitled to receive profits. Okay. Minor, can he be a partner? Minor cannot be a partner, but minor can be admitted as a beneficiary. But how long he can be a beneficiary? Until he attains majority or Whenever he gets to know that he has taken as a beneficiary. So 18 or whenever I get to know I'm a beneficiary, whichever is later. So that means I got to know when I was 30-year-old. Until that time beneficiary only, huh? Whichever is later, no? 18 years or whenever I get to know, whichever is later, I got to know when I was 30. Until then I'm a beneficiary, huh? The maximum time given to you is 6 months from the date of majority. You can't take your own sweet time. Maximum limit is 6 months. Sir, within 6 months also I do not communicate my decision. Then what will happen? By default, I continue to be a partner. Sir, what if on the 6th month, I will say I do not want to continue as a partner. First of all, from 18 years to 18 years, 6 months, this period, will I be treated as a partner or a beneficiary? Until you give your decision, public decision, until the day, you will be treated as a beneficiary only. Sir, if I am saying I am a partner, I was admitted as a beneficiary when I was 16-year-old. Now I'm giving after 18, I'm telling you, yes, I want to continue as a partner. When will my rights and liabilities start from as a partner? From the day I give decision? From the date of public notice? From the date of 18? Then the day he was admitted as a partner to the partnership firm. That is, people. One place I told you yesterday, there is one exception. When we are doing minor agreement, I told you. Minor agreements cannot be ratified. I told you one exception is there. That is partnership. You will be treated as a partner. You will be liable for all the contracts that the partnership firm entered from the day you were a beneficiary. So from 16 years only you are liable. That's the only exception to ratification. Remember that. Hello. Clear? Yes or no? Okay. Okay. Legal consequences of partners coming in and going out. Admission of a partner. When will his liability start from the? From the day he is admitted to the partnership firm. For the past debts, am I liable? Answer is no. But can I be liable? How? Word, provision. Novation, very good. Novation, the partner can be liable. Yes, correct. Yes, novation, the new partner can be liable. Yes, who and all should agree for novation to happen? A and B are the other partners. C is the new partner. D is the creditor. Who and all should agree? A also should agree. B also should agree. Creditor should also agree. C should also agree. Everyone should agree. That's when the novation will come into picture. Agreed? Sir, A left the partnership firm and went. After leaving the partnership firm, is A still liable for the old debts? Think and answer. Okay, A left the firm on 1st Jan 2020. 1st Jan 2026, he left. Public notice was also given. But there was a contract we entered on 1st Jan 2025. We had taken a loan. For that loan, after leaving the firm, after giving public notice also, is A liable after 1st Jan 2026?
No, sir, he's not there.
Is he liable
No, sir.
after public notice?
He's not there.
Pramod, tell them.
He's not liable.
He's not liable. Why? Da?
Because he gave public notice.
Because he gave public notice.
Like he's liable.
A is liable, people. Public notice, once you give, you're not liable for new notices, new contracts, new agreements. Future, you are not liable. Past, Katham, you are liable. What does it say? See here. Pramod, with consent, agreement, one can retire from the firm. His meaning what? If at all something happens after me giving a public notice, if a new loan is given, then for that I will not be liable. But whatever happened, because what happens, people? See here. Understood? Huh? Hey, what is with this subject to novation done? Now A, B, A, C, A. D gave the loan. Agreed? Huh? Who is leaving the firm? A, na? Macha, go and ask B. I will go out of the firm. Please exclude me from the past liabilities. Please. B agreed. I'm going out of the firm. Please exclude. Agreed. Agreed. There is no. Someone said something? Yeah, wrong. Okay. So B, C, and D, all of them agreed. Now in this case, novation. Can I now be excluded from the liability? Answer is yes. Again, parties to the contract are changing. Yesterday only I told you, if at all for the same agreement, the names of the parties change. It is always called a novation, not an alteration. In Indian contract also you saw what are the contracts which are discharged. When are the parties discharged? Now A can never be held liable because you have discharged. Hello? Agreed? Huh? I don't know how much you guys are understanding. Understood, Ada? Okay, good. Taka will finish it off, huh? Indian partnership, maximum another 10 minutes. Tell me now, how do we plan? What do you guys, luncha, gincha, yeno? If lunch, tell me time now only. That's the time. If 12:30 can work, we can finish this chapter. You guys can go for lunch and come. Or if you're okay, then no, we'll finish this unit. After that, you will go for a break. You will come back and then we'll continue. Or if you want, so 12:30 you will take a break. 12:30, 12:40. Yes. Companies Act, promise on you, I'll finish. 100% today only. Maximum I'll take for entire Companies Act. Let us imagine 1 hour. We'll finish it. Negotiable instruments, another 1 hour. So let us imagine even if you go by 12:30, if you come back by 1:30, 1:30 to 2:30 Companies Act. Negotiable instruments, another probably say worst case 45 minutes. 2:15. LLP 20 minutes. So let us add another half an hour to it. 3:30. Yes, we are in a good shape. We can finish it. 2 o'clock. Lunch. ಅದನ್ನ ಹೇಳಿದ್ದೀನಲ್ಲ ಹೇಳ್ತೀನಿ ಚೆನ್ನ ಹೇಳ್ತೀವಿ ಓಕೆ ಫಸ್ಟ್ ಇದು ಮಾಡೋಣ ಅಲ್ಲ ಫಸ್ಟ್ ವಿಲ್ ಡೂ ಆಮೇಲೆ ವಿಲ್ ಫೈಟ್ ಎಸ್ we'll fight for some time. We'll finish this unit and fight down. We'll finish Companies Act also. Okay, easy unit, Sina. Nothing is there. Yes, 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 yes. Hello, the distracted crowd. Not right. ಆಯ್ತಾ huh? Expulsion we did not do. Oh my god. Expulsion of partner. Hey, what do you mean expulsion of a partner? Da? Huh? Expulsion of a partner is nothing but people removing a partner from a partnership firm. Can we remove a partner? Provided it should be in the interest of the partnership firm, not for your personal benefit. If that is the case, yes, removal is valid. So for the removal to be valid, people, certain things has to be satisfied. What is that? First one, power to remove a partner should be there in the agreement. Next one, majority of the partners should have voted for the removal. It should not be one person's decision. And it should have been exercised in good faith. Remember, you can expect a question here. Good faith means what? You are removing him for a genuine reason, not your personal agenda. You have some personal conflict. That's why you want to remove that person. That cannot be a reason for removal. If all these three conditions are satisfied, then removal is valid. If not, removal is considered as invalid. Now, good faith means what? Expulsion to be in the interest of partnership, not your personal interest. For the purpose of partnership, you remove him. It's okay. A notice of removal to be served to the partner. Last one, opportunity of being heard. What is this? Principle of natural justice. Before hanging him, ask him, is it okay to hang you? Son. If you say no, we'll again hang him. Such expulsion is null and void. You remember yesterday I told you, beyond Supreme Court also, if at all there is a death sentence passed, hanging, you will have one final option. You can write a letter to President of India. If Supreme Court also says death penalty, you can still try your luck. President of India, please excuse me. For example, Ajmal Kasab wrote a letter to President of India, your Mumbai attack. Supreme Court has passed death sentence. It was finalized that he will be hanged. So he wrote a letter, dear President of India. When was it? I'm saying you are applying. I'm not saying he will approve. You will file an application. That's all. That's the perspective I'm saying. Now, people, so I'll file it with the President of India. Now, Ajmal Kasab filed. Please excuse me. By mistake, in some state of mind, I just killed some 100 people. So please excuse me. Did we Papa da, he's died. It's passed away. He was executed. The plea was rejected. But I'm saying, yes, it is possible. In, I think if I'm not wrong, this place I might not be very 100% sure. 2005 or 2000, Allah Guru, this is different. 2005 or 2015, that was the first time where we have executed one woman for the first time, one lady, serial killer. I think it was in the year 2005, if I'm not wrong. Yaar nangu gottilla. I forgot name and all. That's the first time that happened. India. She was a serial killer. She had killed children. Kids. How many people are that? I vaguely remember this was there when I was doing LLB. It's been a long time, so I don't remember accurately. But that was a time where first time the lady, one lady was executed. Okay. Next one is people, insolvency of a partner. What is insolvency done? From the day a partner becomes insolvent, from that day, his assets are no longer liable. For the previous acts, the insolvent partner's assets will be liable. From the day he is declared as an insolvent, from that day his assets are no longer liable. Liability of estate of deceased partner, what do I mean by that? Deceased partner means a person who has passed away. The day of death, from that day, all your assets will cease to be the part of partnership assets. Any new losses, any new obligations, your assets are not liable. Past, liable. Your assets are liable, but for the past, but not for the future. From the date of death, from the date of insolvency, your liabilities come to an end. Remember, exam, they've asked you a question in this part. From when will it come to an end? Hello? Clear? How many people have been hanged till now? I'll count and tell. Hey, hey, you're all used to so much used to chat GPT. Correct, Oda? Partnership firm. Pramod? All good now. Yes, here. Partnership firm. Okay, last chapter, last unit, here. Now, people, if at all, registration of partnership firm. Now, whenever is partnership firm registration, is it mandatory? Registration of partnership firm, is it mandatory? Answer is no, it is optional. But remember, even though we say it's optional, you will not enjoy any benefits if you are unregistered partnership firm. So indirectly, you are compelled to register. Today's date, though, you don't even have a choice. For example, imagine you are a partnership firm. You want to sell something on Amazon. You want to sell something on Swiggy. You are a probably say a hotel business. You cannot do it if you are not registered. These platforms will not accept you without certificate of registration. That's what I'm saying. When the act was made, yes. But today's date, all this small, okay. Simply say, yes, it is optional. But in real life, it cannot exist at all. Clear, huh? But yes, as per the book, it is optional. We give all the necessary information to a person called as registrar of firms of that particular area. If whatever information you guys have given, if it's fair, fine, true, accurate, the registrar will give you a certificate of registration, that is incorporation. And remember, there can be a scenario. A partnership firm was registered in, it was set up in 1990, but they want to register it today. Is it possible? Yes. Just that you need to pay something called as late fee. Because you were set up in 1990, in 2020, now it is 2025. What were you doing? So for that, you have to make good. For each year, you need to pay 100 rupees. So if it is 35 years, you need to pay 35 into 100 rupees. That's a late fees. Can you still register? Answer is yes. One question that they could have asked, but they have not asked till now. You know what is that? If a partnership firm is not registered, can I file a case on the third parties? Is it possible? But third party can file a case on you. Now let us imagine there is a case, the partnership firm is not registered and the event happened. Whatever, imagine we had to get money from them, they have not given us. We are unregistered partnership firm. Can I get registered now and then file a case on them? Subsequently, can I get registered and then file a case? Possible? Possible or not possible? Logically think an answer. When the event happened, I am unregistered. Can I later register and then file a case? Pramod, what do you think? Thinking. Huh? Possible? The left hand side. Possible, not possible. Not possible? Of course, how can it be possible? Correct, no? Possible, not possible. Possible, not possible. Possible. When should you register is not given.
When you want to file a case, you should be registered. That's all. You can subsequently register and then file a case. Allowed. Understood? What are the disadvantages of non-registration? One is you cannot file a case on third parties.
No set off.
You cannot claim set off. What do you mean by set off? Sir, we had given them some money, sir. They had given us 1 lakh. We have also given them 20,000. They can't set off that money. Imagine if they have given us 1 lakh. We have given them 20,000. Technically, how much we should pay? 80,000. But they have filed a case on us for the entire 1 lakh. We cannot tell in the court, sir, we have paid them 20,000. I get the point. Pradeep started saying, sir, it's unfair. How fair is it? We have paid 20,000 and still they are claiming 1 lakh. It's unfair. Pradeep literally started crying there. Now, because Pradeep started crying, they made a law. What? We will allow you to set off, but not more than 100 rupees. Now we'll ask, Pradeep, are you okay? Are you happy? Are you satisfied? Now, how much you paid? 1 lakh. I will allow you to set off 100 rupees. Now, just to pay 99,900. Okay, na? Happy or not? Yes or no? So, people, remember, even if you are unregistered, you can claim set off, but not for more than rupees 100. Understood? Yes, sir. 1872, that time it was made. Oh, sorry, 1872 only. Indian Partnership Act was also part of Indian Contract Act only. In 1932, it was separated. So the word 100 was written that time only. Clear? Hello. Aggrieved partner cannot bring legal action against the firm or partners, but he may go for dissolution. Meaning, one partner did fraud. We cannot go and file a case on him. But sir, I don't want to continue with these partners, sir. Please give us dissolution order. I will go home at least. That is allowed. But amongst you, you cannot fight. Let us imagine there is a death. A legal representative did not get the assets of the partner. He wants to go and file a case on the unregistered partnership firm because he did not get his settlement. Can he go and file a case? Answer is yes. A, B, C. C died. C's legal representative did not get the assets, his share. He wants to go and file a case on this partnership firm. Can he file? If you are unregistered?
Yes. Yes.
Answer is yes. Third party can sue the firm. Exception, non-registration of partnership does not take away these rights. What? Third parties can sue, partners can sue for dissolution or settlement of accounts. Here they can ask you a question. Power of assignee of court to release property of insolvent partner. What do you mean by that? ABC is an unregistered partnership firm. C became insolvent. Court appoint a liquidator to come and take the possessions of C's property. Now, can liquidator come and file a case on them, or can liquidator come and sell the property of these particular partnership firm? Whether you're registered or unregistered, if the court is appointing a person, yes, you have every right. Next one, you can claim set off up to 100 sued by legal representative of deceased partner to realize property of the firm. Exam, you can expect a question here. Remember and go. Next one, effect of change in constitution. What is that? Remember, people, in short, A, B, C. If a new partner comes in, earlier A, B, and C was registered. A new partner came in. It is your duty to intimate this as well. If you do not intimate an addition of a new partner, you will be treated as an unregistered partnership firm only. Every addition is also considered as a reconstitution. If you do not communicate it, you will be considered as an unregistered partnership firm. So if you want to file any case after a new partner has joined, it is your duty to first register and then file a case. Sir, but whereas, let us imagine there are
A, B, and C are the partners. C passed away. We have not yet intimated to the registrar. Only A and B are continuing. We did not intimate about the C's leaving us. Now, is this considered as a registered partnership or unregistered partnership? You will still be considered as registered partnership only. Why? In the registrar's books, A's name is also there, B's name is also there. There is no new party that has joined. You will be still given the same benefits or rights of the registered partnership firm. Whereas in the previous case, A, B, C, D, D's name is not there in the register of the partners, whichever is maintained by the registrar. He does not know about D. That's why we consider it as unregistered partnership firm. If you are a partner, we should know. If you are a partner and if it is not communicated, I will treat you as an unregistered partnership firm. Because end of the day, what do you mean by firm? Partners collectively are called as firm. If I have to call only A, I will call A, come here. If I have to call B, I'll say B, come here. If I have to call all four, A, B, C, D, come here, I'll say firm, come here. Firm is not an artificial entity. Four people put together collectively is called as firm. Now, according to A, B, C, and D, they are four. But according to registrar, only A, B, and C are called as firm because we do not know about D. That's why we are treating when a new partner is coming in. I'm treating you as an unregistered partnership firm. His name is not included. Hello?
Yes, sir.
That's the logic. Understood, huh? Okay. Next one, sir. Modes of dissolution of firm. Voluntary dissolution. Next one, sir. Dissolution of firm. How and all can a partnership firm dissolved? One is voluntarily. One is by the court's order. Voluntarily how? Dissolution by agreement. One is follow whatever is there in your agreement. According to that, dissolve. Next one, compulsory dissolution. When will this happen? All the partners will become insolvent. Or there are 5 partners, 4 become insolvent. One person, what will he do? Everything is considered as, again, dissolution. Happening of event which makes it unlawful. What do I mean by that? ITC company, imagine, if it is a partnership firm, if they're doing only pufu, court passes an order. Going forward, in India, tobacco is illegal. And I'm doing only one business. What else I can do? I have to dissolve the partnership firm. Agreed or not? Happening of contingencies, meaning we clearly told upon this event, we will dissolve. Example, partnership for fixed period, 5 years. We said we will dissolve. After 5 years, you have an option. If you want, you can dissolve. If not, if you want, you can continue. It is completely your discretion. If you continue beyond that 5 years also, it will be called as partnership at will. Correct? Huh? Completion of the specific business, metro completed, you will dissolve. Death of a partner, remember, this is optional. If A, B, and C are there, if A, B wants to continue, they can continue. But what if A and B alone are there? B dies, it will come to an end. Adjudication of partner as an insolvent. Same thing. If partners become insolvent, it will be considered as dissolution. Dissolution by notice of partnership at will. At will means when? By if any one partner decides we have to dissolve, we will dissolve. What will be the effective date of dissolution? If at all the partner has clearly said from 1st Jan 2026, the partnership firm stands dissolved. If the date is mentioned, then it will be from that day. Sir, if the date is not mentioned, then from the day the communication is given, meaning I informed everyone on say 10th of December, from that day it will be considered as date of dissolution. Clear?
Yes, sir.
Next one, sir. Dissolution by order of the court. When? First one, whenever a partner becomes insane or unsound mind. But remember, this will not apply for a sleeping partner. We are only saying from the active partner point of view. If a person becomes an unsound mind or an insane person, the other partners or the partner's relatives, they can apply for dissolution. And if the court is satisfied, then only they will order for dissolution.
Remember, temporary sickness is not one of the reason. It should be permanent sickness. Yes, sir. Permanent incapacity, strawberry juice. Active partner is no longer able to work. Can be a brutal accident. That is called as permanent incapacity. Hello? Misconduct. What is misconduct? Misconduct. Illegal activity is misconduct. Anyone in the recent time. Okay, let us imagine the A, B, and Vijay Mallya are the partners. Will you guys do business with this partnership firm? Why? Huh? I'm asking, I'm saying, I did not say you should not do. I gave you guys a choice. Will you guys do a business with him? Huh? Court won't allow? Well, what if you go and do it in UK? Podcast only they allowed. Yes, sir. The people. See, because if he was in India, if which celebrity can come and speak about a case that is going on in the court? Because you cannot speak. Whenever there is a proceedings, legal proceedings, you are not supposed to speak. This he did not speak publicly. He spoke in the room only. That's okay. Sorry. Correct. That's why, because the rules of the country did not apply there. He followed that country law. Yes, no? Okay. Now tell me, you will do the business, Anna will do. Okay, you will do, Okay, you will not do. You have your own opinions, Now A and B are feeling, Macha Vijay Mallya, because of you, we are getting affected. Because of you, we are getting affected. If you can prove it, then people, that can be one of the reasons. He has not done anything illegal. We don't know. But is it affecting the business? Answer is yes. Hello? Okay. That is only called as what? Misconduct. It can be in his personal life or in the business. Anywhere. If it is affecting the business, yes, I have a right. Breach of agreement relating to management of affairs. Embezzlement means what? You're taking money illegally. Erroneous accounts, you spend 100, but you say it as 1,000. Holding more cash than allowed. In businesses, generally, there will be no cash transactions allowed beyond a point. For example, I keep saying that. Now, for example, most of you have done admission with Arivu. Yes. Some people have done with Arivu. How many of you have paid money in cash? I'll say 4 branches. The cash transaction will be. You prove me wrong. Yes, by mistake also there will not be even one admission in 7 years in cash. We pay outrightly whatever is the GST required for the government. Now I'll tell you, I don't know, have you guys been in different places? Have you given cash? I'll not even tell you. Anyone is taking cash, trust me, they're beating the system. Anyone. Cash today is nothing but, I do not want to show the account of it. Now, for example, don't you think, now we do not take salaries in cash. Everything is bank transfer. Everything, every rupee. We all pay our IT returns. Because we are coming and teaching you law. And imagine in the background, if we don't follow law, can we keep our chin high and can we speak about it? Answer is no. And that confident we are. Even by mistake, even one employee wouldn't have compromised and said, it's okay, sir, you give in cash. 500%. No matter where you go, that is the rule. Yes, say something about the system, right? Yes, good. Will it come with the cost? Yes. We will pay GST, higher rates, yes. But that's how the system is, right? If everyone starts thinking with it, then how will the country prosper? Yes, no. So some good is good. Okay, transfer of interest to third party. A and B and C. Remember previous example. C asked A, Macha, please buy my share. A said, no, I don't have money. B, you should buy. I don't have money. Hey, D, you at least buy da. D purchased, outsider. Now he came into the business. A and B does not like D. Now people, what they have a right. They can come and apply for dissolution. Sir, we do not want to continue. Please allow us for dissolution. Exam, they can ask you a question. Sir, is it a mandatory? Yeah. Look at the words. Continuous or perpetual losses. Just an equitable grounds. A discretion of partner. What is this? The just an equitable grounds. The hey, this continuous or perpetual losses. Remember, I think once they have asked the question, A, B, C, they have incorporated a partnership firm registered for 5 years. For the last 3 years, only losses. One of the partner is of an opinion that we have to wind up the partnership firm. A and B says, no, we have to continue. They'll ask you, does C has any option in this given case? Can C do anything? C can apply for the court for dissolution under the grounds of continuous or perpetual losses. Understood? Huh? When will we come? Generally, students will ask, sir, why can't you go voluntarily? Now, A and B does not want to dissolve, but C wants to dissolve. When you guys cannot act together is when you will come and seek the court's route. When you're acting together, easiest. Agreed? Huh? Next one, just an equitable. Just an equitable is nothing but people, etc. I can't write everything. Da. So one of that is deadlock of management. Deadlock of management means what? We have 4 partners. 2 says yes, 2 says no. What to do? It's called deadlock. They are not able to convince them. Then what? How do we go forward? They are not able to go forward. Then that's all dissolve. Next one, management not in talkative terms. Fight on, in and out. I'll not like you, you will not like me. It'll continue. How will the business go on? The third one, loss of substratum. What is the substratum? We started for a particular purpose, or we started for a particular object. Now that object is no longer prevalent in our society. For example, we started typewriters. Can we still keep doing typewriters? If you are updating yourself, okay. If not, loss of purpose. Meaning, we also call as obsolete. Obsolete means people, the product goes away from the trend. Such products are called as obsolete. Yes, sir. Loss of substratum. The purpose is no longer achieved. Agreed? Next one, gambling by partner on stock exchange. One partner takes all money. He said, I will double it. He doubled it. 3 zeros were there. He doubled it this side also. Yes, sir. So people, this is called as gambling by partner. Again, one of the ground for dissolution. Then, just one thing that is there, what dissolution of firm and dissolution of partnership, are they same? What do you mean by dissolution of firm? End of the partnership firm. Dissolution of partnership. A, B, C is going out. It is a dissolution. D is coming in. Dissolution. So here reconstitution happens. Here liquidation happens. Here it will be realizing of assets. In reconstitution of firm. In reconstitution of partnership, revaluation happens. Reconstitution of firm, the business will continue or business will come to an end. Business will continue in the case of partnership or dissolution of firm, dissolution of partnership. Dissolution of partnership, it may continue. Dissolution of firm, business will not continue. Agreed? Dissolution of partnership may or may not lead to dissolution of firm.
But dissolution of firm will definitely lead to dissolution of partnership. So go for a break and come. What time we are catching up? 1:30? 1:40? Okay, 1:45. 1:45, okay?
No, I will, Papa, inform the next faculty at least. Mentally, you should be correctly in correct state. Okay. No, you're all. No, hey, online, I didn't tell you, da. Not you, I said to them. All of you are brilliant, simply I said, huh? Yes or no? No. See how fresh and beautiful and you guys are full. Sir, yes, sir. Yes, sir. Next topic. We know this. Go to next topic. That's how you are. See, enthusiastic souls. Okay. What plan tomorrow? Sleep. I thought of having class at 7. 7? 7 is okay, no, da? 7 is okay, no? 8 is okay? Okay, God's grace depends on your friends and cooperation. Okay, no one is there, no? Okay, so if you guys are finishing it today, we'll finish it today. Tomorrow take a day off. Yes, sir. So let us start the Companies Act. Easiest chapter of all. Yes or no? Direct question, no? There will be little indirect questions also, but no and go. Very, very important. So let us start our next chapter, sir. Companies Act. Yes, people, tell me, what is company? Tell that clearly. What is a company? అవును ముందుకు నేను యూజువల్లీ టెల్ ఎస్ ఎనీ అదర్ లా ఐ హర్డ్ ఇస్ ఓ సారీ డా మై మిస్టేక్ okay company means what people company means a company registered under Companies Act or any Companies Act 2013 or any other previous company law that existed. So any other previous law. Such things are called as what? Companies. What are the characteristics of companies? Separate legal entity. What do you mean by that? Company is different from members. Then why are we behind Vijay Mallya? Lifting of corporate wheel? What do you mean by that? Members are treated as different from ಅರ್ಧ ನೀವು ಹೇಳ್ತೀರಾ ಹಾಫ್ ಐ ವಿಲ್ ಟೆಲ್ members are distinct from the company. Okay, fair enough. Now people, characteristics of a company, yes, as you guys rightly said, what? There is something called as separate legal entity. That's the nature of a company. Separate legal entity means what? Company is different and members are different. In short, what do you exactly mean by this? Now, for example, who is the founder of Arivu? Arjun sir. Now Arjun sir wants to see India South Africa match, which Indians are playing really good. So we want to watch it in a bigger screen. So Arjun sir wants to take this TV to his home. Can he take it? Why? So people, even though the company belongs to a founder, the founder himself cannot have even one asset belonging to the company with the founder. Not possible. Now this concept is called as what? Separate legal entity. My assets are mine. The company assets belong to company. Whereas in partnership, that was the difference, isn't it? We said, right, firm means what? All the four partners together, I will address it as firm. That's all. Partners are not different. Partnership firm is not different. They are all one and the same. Together we are addressing. See, I can't call A come, B come, C come. I'll say A firm come. But when I'm calling in the other case, if I'm calling a company, I'm not calling the shareholders. Company will be liable. For example, Byju's. Now it is going on your insolvency and all of that is happening. There's so much of debt to repay. Now are the founders responsible to repay that? It's a business loss. The founders' assets are safe. You will not question the founders' assets. Dream11, Paytm, what and all, Videocon, so many insolvency cases are happening in in India. For all of that, we will not ask the shareholders to pay from their pockets. I mean, I would have told this to you in the class. There was a company called as Videocon. Videocon, there is a, liability for Videocon. What is the liability of Videocon? The liability of Videocon was around 74,000 crores. That's the total liability of Videocon. How much assets they have? Around 2,500 crore. But we are not touching the founders. You guys don't even know the founders' names. But we know Vijay Mallya. Papa, 6,000, Papa. Inhuman people. 6,000 crore, you guys made his life so miserable. Where is 6,000? Where is 74,000? Hello? Then? Because Videocon failed as a business decision, not because of manipulation or misappropriation. Genuinely, if a business fails, we will not ask the founders to pay the money, or the directors to pay the money, or the shareholders to pay the money. The company's liability is companies, the shareholders' liabilities are shareholders. Both cannot intersect. That is theirs, it is theirs. Whereas in partnership, that was the risk. If anything partnership firm does, unlimited liability, right? You are liable. If partnership firms' assets are not sufficient, money will be taken from your personal accounts. Agreed, huh? That's what is called as people separate legal entity. The case law also you would have seen something called as Salomon versus Salomon. Again, I'll put it in the case law only. Let us see that in there only. Next one is called perpetual succession. What do you mean perpetual succession? Members may come and go. Company will go on for ever and ever. Tata Steel, when was Tata Steel incorporated? 2018? 18th century? 1818? 1880s? So people, Tata Steel, pre-independence companies, they are more than 100-year-old. Formal structure came in 1915, but they existed since 18th century, Tatas. In fact, Tatas are the first people in India to introduce Sundays. But for others, Sunday was introduced because of 1947, 1950. There were so many acts passed. Tata said when people are working for 7 days, let them rest for 1 day. That's how the concept of 6 days and 1 holiday came. Maternity Benefit Act came in 1950s in India as an act where the employer had to pay leave for pregnant women. But Tata's implemented in 1905. Yes, sir. So 19th century, who was the person who, probably registered Tata? Jamshedji Tata, it goes, no? Jamshedji Tata, then comes Ratan Tata. Now Ratan Tata is also no longer there, but Tata is continuing. Yes. Did Tata take an effect because of it? No. Members may come and go. Jamshedji Tata, Ratan Tata, but the company will go on forever. Company's existence, did it come to an end? No. It is still continuing. Yes, sir. That is what is the meaning of perpetual succession. Nominees, legal heirs, they will continue. Another example, Reliance. Who started it? Dhirubhai Ambani. Who is running it? Another person also is there, Papa. Yeah. Anant Ambani. Okay, limited liability. What do you mean limited liability? Correct? Liability is limited. To the extent of your whatever is my capital, to that extent I am liable. Artificial legal person, the company can enter into contract in its own name. If you have a problem, you will file a case on the company and the company can file a case on you as the case may be. So in India, in the eyes of the law, we consider company as another person, just like you and me. Next one is common seal. What is common seal? Signature of the company. So if company wants to enter into a contract, how will they enter? They will say on behalf of the company, if you affix a common seal, that is sufficient. But remember, today common seal is not mandatory, common seal is optional. In 2015, they passed a amendment. They said, why the common seal is mandatory? You only logically think. What are we telling? If company wants to enter into a contract, we are telling you have to affix a common seal. Common seal, who is affixing? What? Company only will come and press the seal? No, one human has to come and press it. Instead of him coming and pressing the seal, can't I just tell you, instead of affixing the seal, just to sign it? Both are same only, no? You can at least save some 1,500 rupees. That is what they said. And that realization came in the year 2015. So in 2013 is when they said the common seal is optional. Sir, so someone has to come and sign. No, who will have to come and sign? They said the alternative is 2 directors will sign or 1 director and 1 CS will sign if appointed. If a CS is not there, then it will be 2 directors only. You can expect a question here. Remember and go. Case laws, okay. Lifting of corporate wheeler. Correct, huh? What is lifting of corporate wheeler? Members. So generally what do they say? There is a shareholders, there are shareholders here, there is company here. In between them people, there is always one line separating them. Agreed? For whatever happens on the company side, shareholders will not be liable. Whatever happens to the shareholders, company will not be liable. But people, if something happens to the company, the liability of the shareholders is always limited. But people at occasional cases, some cases, they will say for whatever is a liability that the company incurs, for that liability, the shareholder will be liable, and that concept only we call as lifting of corporate wheel. The curtain in between them, the separation in between them will be lifted and the vertical lines will become horizontal lines. Whatever is the act done by the company, the shareholders will be responsible. Whatever Kingfisher did, there was some part of it as a guarantor that the Vijay Mallya was affected, as a director, as a shareholder, for certain decisions he took, he was affected. The decisions was like misappropriation of funds. He suggested, see, if you look at that podcast, in that he said it was a marketing campaign. But they said, people, marketing is fine, but you spent way too much of money on Formula 1, Royal Challengers. But why did we give the loan? Banks said, why did we give the loan? We gave the loan for Kingfisher Airlines to operate. But you spent that money on these places. So they said you have misappropriated the funds. On that capacity also you are liable. And that's why we are behind Vijay Mallya for so many things. Understood? Yes, sir. So what do you mean by lifting of corporate veil? Generally, the liability is limited. But people, in occasional cases, whatever actions done by the company, if at all it is not right, if it is illegal, in that cases, people, we will say the limited liability will come to an end, the shareholders liability will start, and that is what is called as unlimited liability. Correct? Sir, when will we lift the corporate wheel? When will we say that for whatever company did, the shareholders will be liable? When is that? One scenario, people, is called trading with alien enemy. When did this happen, sir? Trading with alien enemy. Trading with alien enemy, people. What is the scenario? there was one company people which was registered in UK. There was one more company people in UK only. Now, the company A was selling some, tires to company B. There was a contract between A and B that we will supply the tires to you, you can sell it. Now, what did company B do? After a certain time, 6 to 7 months, company B said, we do not want to purchase the tires from you going forward. Company A said, that's a breach of contract, we will file a case on you. Company B said, even if that is the case, we will still not buy the tires from you. The people, there was a dispute. Company A went to the court, filed a case on company B. So there was a contract that they have to buy the tires from us for 5 years. But after 6 months, they are telling we do not want tires. So we need compensation. Company B was asked, why did you guys want to stop this contract from company A? What is the reason? They said, sir, because company A is our alien enemy. How can they be your alien enemy? You are also in UK, they are also in UK. How can you both be alien enemies? They said, people, the company A, who are the shareholders of company A? The shareholders of company A people were from Germany. They were all German citizens. They had started the company in UK. Now, when this entire case was going on, there was World War going on. UK and German had treated each other as alien enemies. They had declared each other as alien enemies. Now, company A said, sir, yes, that is correct. We are alien enemies. But, sir, there is a separate legal entity. No, sir, my shareholders are there, but I am here. So, whatever we do, they are not liable. Whatever they do, we are not liable. There is a separate legal entity concept. We are different from our members. But people in this company B said, sir, okay, let us assume what they said is correct. Let us imagine we go ahead with this contract. We give them good money. Sir, they earn good profits. Yes, correct. If their profits goes up, their dividends will be declared. If dividends are declared, don't you think, sir, we are indirectly giving money to our alien enemies only, and we are the reason for it. The court said, yes, whatever you said makes sense, sir. Corporate wheel was lifted, and in this case, it was decided, people, whatever are the actions done by company B, stopping of the contract was considered as valid. Why? Corporate wheel was lifted, and it was came to the light that company A and its shareholders are one and the same. Lifting of corporate wheel. Understood? Hello. Why did we lift? To figure out what? Whether are we entering into a contract with a alien enemy. Case law, Daimler Company Limited versus Continental Tires and Rubber Company. Clear? Hello? To evade tax, what happened? One day, there was one person, Anna had good income. What did Anna do? Anna formed 3 dummy companies, company A, company B, company C. He had 1 crore rupees. He split that money into 40 lakh, 30 lakh, 30 lakh. What did these companies further do? These companies further invested in other companies like ITC, Tata's, Reliance, Infosys, more companies. They further invested. Now, of course, when imagine you invested in ITC, you invested in Reliance, they will start giving you dividends because their performance is good. Agreed? Now, company A started earning profits. Company B started earning profits. C, profits. According to Income Tax Act, whether you earn money or company earn money, you have to pay tax, no? Now, company earned money. Should they pay tax on it? Answer is yes. Now, what did this person do? Person sitting on the top. He borrowed money from these companies further. Imagine company A earned 1 lakh rupees as a dividend. What did company A do? Company A gave this 1 lakh rupees to this person as loan. Company B, whatever they earned, they gave this money to this person as loan. Company C, whatever they earned, they gave that money to this person as loan. Of course, end of the day, the entire company belongs to him. He never repaid those loans back. Now, there were profits, but they gave loans which never came back, which became bad debts. Technically, what happened? Company A, company B, company C, none of it paid income tax because everything was bad debts. Okay, now this person took money from the companies. No, should he pay tax? Why will he pay tax? In which country you will pay tax on loans? So in this way, what did this Anna do? He literally evaded tax for almost like what 6 to 7 years. Again, what did we do? Lifted the corporate wheel. They said the company A, B, C, and this person in the top. They are all one and the same. The case law, Dinsha Manekji Petit's case. I didn't get you. Little different. Ponzi schemes are nothing but a scheme which is not registered any other place. This is nothing but manipulating the system. Ponzi scheme, if I have to give you a perfect example, network marketing, your word, I will join you. You join another 10 people. You heard, that is only called as Ponzi scheme. Yes, clear, hello? Case law, Dinsha Manekji Petit case. Okay. Third one, subsidiary to act as an agent. What happened in this case? There was a company who was into logistics transport business. They applied for some licenses for their vehicles with the British Transport Commission. Because they did not comply with certain laws, British Transport Commission rejected their license. What did this company do? This company formed one subsidiary company. They again applied for license. Their idea was, if we only apply, our application will definitely be rejected. Because they rejected the license saying that you have not completed all of this and you cannot apply for a license again for a certain period. So what did they do? They formed a subsidiary company. Through that they again applied for a license. Now British Transport Commission figured out people. They said this company and this company are one and the same. This company is trying to do something indirectly. They could not do. That's why they are doing it indirectly. And British Transport Commission rejected their application also, lifting the corporate wheel. Holding company has appointed a subsidiary company. They have formed a subsidiary company to act as an agent. Whatever in their name they could not do, they wanted to do it in subsidiary company's name. Hello. If you guys remember agents chapter, there I told you, undisclosed principal. The third party gets to know who the principal is. They can revoke the contract if the contract is not yet completed. You remember, Vijay Mala example I had given you there also. Loan. Okay, that is the case, people. Merchandise Transport Limited versus British Transport Commission. People, same cases will be asked in your exam. Same stories will come. Hello? Okay, next one. To avoid legal obligation. What do you mean to avoid legal obligation? One day what happened? There was one company, company A. Company A had good employees. According to the law of the land, what is the law? Whenever a company earns good profits, that means it is because of employees' effort. So they will have to give bonus to the employees. That was the rule. Now people, as the days passed by, company A earned good profits, their bonus also went up. In addition to that, company A had some investments in another company. They had extra money, no? They've invested some money in other company. They made investments. Now, of course, they also started giving dividends or interest, as the case may be. Again, people, company A's profits started going up, because of which bonus also went up. Now, what did company A think of? Hey, why are we giving them so much of easy money? Let us do one thing. Let us take off these investments from our name. They transferred all these investments to the name of company C. They formed one more company called company C. Now, what did company C do? They formed company C. Whatever shares company A had in company B, they transferred everything to company C. Now, company C is a shareholder of company B. Now, when company B declared dividends, now no longer A got it. Because of that, the dividends started going down. Because of that, bonus started going down. Now, they saw 1 year, 2 years. Now, they also suspected something is happening. Now, when they filed the case, it came to the light, people, that company A has done such arrangements to reduce their profits in their name so that they can save the bonus payment to be made to the shareholders. Corporate we lifted, they said company A, company C is one and same. Whatever profits was made by company C, they had to pay certain commission, certain percentage as bonus to the employees. What is that, sir? That is only the case law. What is the case law? Workmen of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. The last one, sir, company formed for fraud. What happened in this? There was a company, Clifford Motor Company. They hired one managing director. That person's name was called as Horn. Now, what was this person's role? He was a MD. When we appointed him, we clearly signed one agreement. Macha, whenever you leave the company for the next 3 years, you are not supposed to do any businesses related to the company. You are not supposed to take our customers. You are not supposed to do anything. Now, what did Horn do? After 6 months, Horn joined the company. After 6 months, the Clifford Motor Company removed Horn. Horn came out. He started selling the spare parts of Clifford Motor Company. Because of which some customers started coming and buying it there. Clifford Motor Company sent a notice to him saying, we clearly had an agreement. You are not supposed to do any business to take our customers for 3 years. So what did Clifford Motor do? What did Horn do? Horn came and he incorporated one company. Who is the shareholder? The shareholders are his wife and his friend. They were the shareholders. But control is with this person. They will listen to whatever he says. I getting the point, huh? Even in our homes also it will happen, huh? Anyone who has gold, property and all clever fathers, they would have all done it in the name of mothers. Anything happens, they will be arrested. Yes, but it is there, no? Why? Same thing, but control. Of course, today it is changing. Today every control is with women only. Yes or no? Yes, sir. Now, people, that is what. Now, what happened here? They opened one company. Now, what did that company started doing? That company started dealing in the spare parts of Clifford Motor Company. Again, people, this time Clifford Motor Company had seen enough. They directly sent a notice to this company. Hey, Horn, how many times did I have to tell you? We told you are not supposed to deal. Why are you doing it again and again? Now, Horn replied saying that the restriction was between me and you. The agreement was between me and you. Company is a separate legal entity. You did not enter into a restriction with the company. It was with me. Horn replied. Now, you tell me, whatever Horn, the company, whatever they did, is it right? Is it right? Now, people remember, as per the agreement, yes, you are trying to play with the artificial separate legal entity. You are trying to play with the character. Corporate wheel was lifted. Who is running the show? It is our Anna. Our Anna is running the show. So, people, the court ordered Horn, you are not supposed to do. Whatever Clifford Motor Company is saying is right. Whatever you could not achieve it in your name, you are trying to do it indirectly. You cannot use the company as a shield to do something indirectly. We will not allow it. And in this case, Clifford Motor Company won. That is the case law, people. Clifford Motor Company versus Horn. Any doubt? Hello? Okay, next one. Class of companies. Different types of companies on the basis of liability. The company can be classified into, first one, company limited by shares. Next one is company limited by guarantee. What do you mean by guaranteed?
The time of winding up, members should contribute to the assets.
Correct. So, on the day one, people, what we give is guarantee. There are two, let us imagine, members. A will tell, I'll give a guarantee up to 50,000. B will tell, I will give a guarantee up to 50,000. The company will start functioning. Now, the company will start to function. Now, people, let us imagine the last day, the company will go on for 7 years. On the last day of winding up, now company will have assets, no? With that assets, people, they will try to repay the liabilities. How much ever we can pay, we will repay. Sir, what if the assets of the company is not sufficient? Now we will come back to and ask, hey, you are told loan of 50,000, come and pay now. Okay, company assets are not sufficient. Yes, company assets completely we have utilized. It is not sufficient. Now people A will come and pay 50,000, B will come and pay 50,000. Such type of companies is called as what people? Company limited by guarantee. They will not give the money on day one. They will give the money on winding up, at the time of winding up, not on the day one. Such type of companies are called as what? Company limited by. In class we would have seen examples. Example, Reliance Foundation is the best example of company limited by guarantee. Reliance Foundation, Neeta Ambani led company. It's a best example of company limited by guarantee. Next one is called unlimited company. What do you mean unlimited company? Simple. The Companies Act has clearly told you the liability of the members is limited. We say no, humko nahi chahiye. We don't want. Why limited liability? I have mast money, I will pay. I said, why da, venda, no, humko chahiye hi chahiye. Now people, law is telling you, enjoy the limited liability. You say no, I want unlimited liability, then die. So simple, it's a characteristic. When you are registering a company, there will be a drop down. You click, it will come as a drop down. You can choose between company limited by share, guarantee and unlimited. You click unlimited, you are unlimited company. That's all. That is how simple it is. The company called as, what do you say? Oh, what is that? Range Rover, Land Rover was an unlimited company till 2013. Later on, they became a limited liability company. Can we change with time? Answer is yes. You can change with time. A company limited by guarantee can become unlimited. Unlimited company can become limited. All that is allowed, possible. Yes, Sam. Pakana. Hello. But remember one thing. The creditors cannot file a case directly on the shareholders. You have to file a case for the recovery of money with the company. Company will recover it from the shareholders and they will settle it with the creditors. Clear? Hello? Any doubts? On the basis of control, companies can be classified into. Company limited by guarantee and unlimited company. Company limited by guarantee and unlimited company can be of two types. First one is called as company limited by shares. Meaning company limited by guarantee having share capital. That is how we call it. Next one is not having share capital. So a company limited by guarantee can have share capital. A company limited by guarantee cannot have share capital also. For example, I'll tell you in simple. I'll give you an example of company not having share capital. Reliance Foundation is a company limited by guarantee. They don't have share capital. Why? They don't need share capital. Why do they need share capital? They don't want capital at all. Why? Reliance Foundation, not Reliance. It's a
Section 8 company.
It's a Section 8 company, but where are they getting money from? Reliance Industries Limited. For them, CSR is applicable. Last year, Reliance Industries ka CSR spend was 1,300 crores. To spend that, they cannot spend it in their name. They will give that money to Reliance Foundation. They will spend that money. Now tell me, why does Reliance Foundation need capital? CSR is applicable. That money is given by Reliance Foundation. Reliance Industries. CSR is nothing. Okay. Corporate social responsibility. Every company earning some good profits you have to spend some money on society. It's a mandatory thing. That is called as CSR. The Reliance Foundation, they'll come and tell, hey, celebrities, give me some funds, da. They won't give, They'll give or not? They'll not give, they played that football match, you remember, Virat Kohli, Dhoni and all. Where did they play? It was a charity raiser for cancer. Who organized it? Neeta Ambani, Reliance Foundation only. Hello? Yes, sir. Why will they not play? Everyone will play. But if one celebrity dances, that will get some views. If every celebrity coming and dancing, money irko. Yes, I need not have to tell you. Wedding videos you guys would have seen. Hey, 3 cans put on same stage, da. And they did dance and all means. Yes, money has value, da. Money plays roles. Correct, Agreed or not? No, people, with this, our Pramod also got inspired. Oh, Section 8 company. Foundation means someone will give money. He also formed Pramod Foundation. Now tell me, will you guys give money or not? No loyalty. CA Foundation. CA Foundation. He will call it as Pramod Foundation. Nitish, you will give it? Nitish only will not give. Why will we go to second bench? Now people, Pramod has no choice. He has to put his capital. That's why company limited by guarantee can be of 2 types. With capital, without capital. People like Pramod will have to put in their money. Not required. He has to put his own money. Yes, sir. At least to start. You have to put no. To become a member, you have to give. Yes. Then how will you become member? What if there is no share capital? How will you become a member? Yes, sir. Hello. Okay. On the basis of control, second type of company is called as what, people? Subsidiary company. How will a company become subsidiary company? Da? Company A. Company A is controlling Company B. In Company B, how many directors are there? 3 directors are there. Company A is deciding who this majority of directors should be. Who is deciding it? Company A is deciding it. So out of 3, 2 directors are appointed or removed by Company A. If one company is dictating that with another company, if one company is controlling more than or majority of the directors of another company, Company A gets the tag of holding, Company B gets the tag of subsidiary. That is the first condition. Understood? Hello. Next one, controls more than 1/2 of the total voting power. What do you mean by that? Company A, Company B, A, B, 51% of paid up equity share capital. Let us assume which share has voting power? Equity. So paid up equity share capital. If Company A is holding Company B, 51% of shares is with Company A. We call Company A as holding Company B as subsidiary. Hello. Sir, there is Company A. There is company, say for example, Company B. Company A holds in Company B 51%. There is Company C. In Company C, Company B holds 30%. Company A holds 25%. What is the role of Company C? What type of company? It's a subsidiary company of Company A. That's the meaning of what? If I hold it, controls more than 1/2 the total voting power, either on its own, everything me only, or together with its subsidiaries. I am holding along with my subsidiary. Together the net is 30 plus 25, no? So it is 55, no? Total in company C, how much are we controlling? Directly I'm controlling 30. Directly I'm controlling 25. Indirectly I'm controlling 30. That means I'm controlling 55. Company C will become subsidiary of company A. Hello? Third option now. Company A, company B, company C. 51%, 51%. This is a subsidiary, this is a holding. This is a subsidiary, this is a holding. This is only called as what people? Deemed subsidiary company. Examples are, this can be what? Walmart, this can be Flipkart, this can be say Myntra. Yes, Myntra is a deemed subsidiary of Walmart. That's how you need to take it. Hello? Done na? Pakka na? Okay, done. There is one more type of company. Company A. Company B. Company A is holding 20%. What is company B? Associate company of company A. What if I am holding 30%? Associate only 30 also. For 30. 40, 50, 50, exactly 50. So remember 20 to 50 is always considered as associate company. Company B is an associate company of company A. Sir, Maruti, sir, Suzuki. There is something called as Maruti Suzuki. This is called as joint venture. Tell me, what type of company joint venture is called? Associate of which company? Maruti Suzuki is associate of Maruti also? Suzuki also? Only Suzuki? Maruti is associate of Suzuki. Suzuki is associate of Maruti Suzuki. Yad Guru is Rangoli. Huh? So remember people, Maruti Suzuki is a joint venture of Maruti and Suzuki. So in the books of Maruti, I will show Maruti Suzuki as my associate company. Suzuki will show in their books as Maruti Suzuki as their associate company. Why? Because the definition says associate company includes a exam question they can ask you. Hello. Pakana. Okay. Next type of company is called as what? Public company. What is a public company? What is the minimum number of shareholders in private company? Private company. Private company. Public company minimum. OPC. What is the maximum members in OPC? Maximum da. Maximum. Maximum. Pramod tell da. When Pramod says it is always right. Now people, what is maximum number of members in private company? When Pramod says it is always public company, what is the maximum number of members? I told you. Unlimited. Agreed? Yes, okay. People, XYZ Limited, ABC Private Limited, XYZ Limited, ABC Private Limited, 51%. Now tell me people, ABC Private Limited, is it a private company or public company? Understood? Private or public? But name as private limited, it's okay. That's okay. Remember people, for functioning purpose, for the functionality purpose, my minimum shareholders, my name and all that, it will be private only. But the role, whatever the rules applicable, for that I will be considered as public company. This is a deemed public company, correct? Cut, copy, paste applies to government company also. A subsidiary of a government company will be deemed to be a government company. Done. Agreed? Next one, type of company, private company. What do you mean by private company, sir? A private company has three things. One is restrictor, next one is limiter, third one is prohibitor. It restricts what? The number of shareholders to what? 200. The maximum number of first restrict transferability of share. In a private company, can the shareholders transfer the shares? You cannot freely transfer. Approvals are required. A, B are the shareholders. Now, if B has to transfer the shares, B has to ask the approval of A. Only then he can transfer. Just like partnership, whatever you saw, same rule will apply. Understood? Huh? Okay. Second one is people limit. What is the maximum limit of shareholders in a private company? 200 members. But when I'm counting 200, I'm not supposed to count a few people. Who are they? I'm not supposed to count. If at all past employees, imagine our employees were there, I've given them some shares. If any employees are given shares, people, you have given them shares, they left the company but they still hold the shares. It's okay, don't count them. Or there are employees who are still with you, you have given them the shares, don't count them. And if there are joint shareholders, meaning what? What do you mean by joint shareholders? Two people holding one share. One share means together they are holding shares. Count them as one and not as two. When you are counting the limit, you are supposed to treat them as one and not as two. Hello? Pakka? Okay, third one, people. There is something called as prohibit. What is prohibit? The company is prohibited from inviting public to subscribe the shares. They cannot go for an IPO. You have to first convert to a public company. Only then you can go for an IPO. It is only private people with whom you can raise money. You cannot go for public. I cannot give advertisement. I cannot give a flyer down. You guys, I'll tell no. Say for example, people, if you guys are interested, you can invest in shares of ArivuPro. We can't do that. Understood all of you? Hello? Next one is called as OPCA. What is OPCA? One person company. Who can start it? A person should satisfy three conditions. What is that? First one, no. He should be a natural person. Next one, Indian citizen. Third one, resident in India or otherwise. If I have to be called as a resident in India, how many days should I satisfy? 120 days in the previous financial year. Correct? Hello? Yes, sir. Okay, sir. In OPC, only one shareholder is there. What if he dies? What will happen? Nominee will come into picture. So should I mandatorily appoint a nominee? Who can be a nominee? Same conditions. A person should be a natural person. A person should be a resident or otherwise, or Indian citizen and Indian citizen. So all three conditions are to be satisfied. Can I withdraw the nominee's name anytime? Can I change the nominee? Can the nominee resign? Everything is possible. You just have to replace the nominee. That's all. Can a nominee be a minor? No. Minor? No. Nominee? No. Not possible. One person can be a member of how many OPCs at the same point of time? Member? Can I be a member of OPC and one private company? Can I be a shareholder of one OPC and shareholder of one private company? Possible? Possible, Possible. Remember, people, OPC there is a limit. You can be a member of maximum one OPC. Private companies, public companies, there is literally no limit. Being a member in OPC, you can also be a member of 10 private companies, 10 public companies. It's absolutely fine. Yes? Hello? Okay. And next, what else? What? Shareholder, what else? In OPC, anything else is there? They cannot convert into a Section 8 company. Can they convert into any other form of business? Can a OPC convert into a private company? Possible? No. Can I convert into a private company? Can I convert into a public company? Is it possible? Yes, possible. Voluntarily you can convert. Absolutely no problem. And remember, OPC cannot carry on certain activities. NBFC, not possible. Non-banking financial companies, I cannot do it. Hello? All of you? Okay. One person can be a member of one OPC, correct? Huh? Simultaneously, can I also be a nominee of another OPC? One OPC, I'm a member. Another OPC, I'm not a member, I'm a nominee. Nominee, da? Nominee, what's the problem? I cannot. Remember, people, one member can be at the same point of time. He can be a member in one OPC, nominee in one OPC at the same point of time. What does the law say? Read. One person can be a member. I can be a member in one OPC, nominee in one OPC. Now your logic is correct, sir. What if wherever I am member, what if he dies? That's why we have second one, no? If at all a member dies, a nominee becomes a member. Now I become member of two OPCs. I have to give away one OPC within 180 days. Hello? Correct? Other type of companies, government company. Government company means what? Correct? Yes, sir. Hello? Now you all know what is government company, no? Pramod? Pakka, no? There is a company called as company LIC. In company LIC, 51% of shares is held by central government. There is a company called company X. LIC holds 15% of shares in X. There is a company X in which state government of Karnataka holds, say for example, 20%. Company X, there is something called Tamil Nadu government holds around 25%. Now they are asking you, what type of company is company X? It's a deemed government company. Why? Jointly you are holding 20 plus 25 plus. Correct, no? Deemed public company. Deemed government company. Hello? Deemed government company. Yes or no? Okay, tell me government company definition. Wait. Central government also let us add. They are also holding 3%. Let us imagine. Okay, we'll come back. In central government is also holding in X. Okay, we'll see. Yes, Pramod, what is the definition of government company? Central government, any state government, or both central and state, or state governments. Again, I am telling you, central government, state government, center and state, or state governments. Okay. Holding together more than 51% of paid up share capital, having voting power. Is called as government company. Now tell me, is it a government company or not? Why is it a government company?
Because all the governments together holding more than 51%.
Where?
20, 25 and
20, 25,
LIC along with the
15. Oh, okay. I forgot this. 15% also you have to take. Again, I'll ask you. Tell me government company definition. Tell me. What is government company? A company which is not less than central government, state government, central and state governments, and subsidiary includes a company which is Oh, includes subsidiary company of a government company. In which place 15% will be called as a subsidiary company?
Central government owns 55% of LIC.
Correct. So LIC is a government company. Okay.
So it is holding 50% of state government.
Now tell me, where is this 15% criteria written in your definition?
Along with the 51,
Where is it written? Show me. Where is it written? Okay, perfect. LIC is considered as deemed government company. Very good. LIC is also government company. You have to add 15% is what you're saying. Where is it written? A provision includes. Tell me, Veda is telling something.
Company which is a
The provision includes.
Which is the subsidiary of a government company also.
Okay, it includes a sub company, a subsidiary of government company also. Correct? Okay, let us imagine there is a company called as Company X. In this, LIC is holding 51%. Now, can I say X is a subsidiary of LIC? In LIC, central government is holding 55%. Now, what type of company is LIC? Government, deemed Allah, government company, because CG is directly holding. Now, what type of company is Company X? Deemed government company. On what provision you said? The provision is simple, macha. If at all a government company, there is another government company, subsidiary of a government company is a deemed subsidiary. Subsidiary of a government company is a deemed subsidiary. This is not subsidiary. 15%, where is it subsidiary? You are not supposed to add. In government company definition, where did they tell you to add this? There are only two cases. Either this, yes, company X is deemed government company. Here you are not supposed to add. So company X is not a government company because the shareholding is what? 45 plus 3, 48. That is not 51%. And hence, this is not a government company. You are not supposed to add this 15. The deemed government company. That is his case. More than 51. Hello. Understood, huh? That's why I told you to say the definition. Where is it written in the definition? Where did they tell you to add this? 15% to be added. Where is it written? Not written, no. Hello? Convinced or illa? Remember the macha exam question, no? Every time we ask, every time it's wrong only. Convinced? So only deemed government company, that is separate. And government company, that's separate. You don't add that 5-10% and all, you're not supposed to add.
Instead of LIC, any private companies, there are also same subsidiary.
Like CG company has invested in A.
Same chart. A private limited. And also 51% in X company.
51%. Same, what difference? You change the name, what else is the difference? A is already a government company, huh?
So A will be holding in extra, it will be a deemed government company, right?
But tell me, where is it written? See, there are only two cases written. A subsidiary company of a government company is deemed subsidiary. For becoming a subsidiary, what is the percentage required? 51%. Now tell me, company X, are they holding 51%? No. Okay, in government company definition, did they tell you to add this case? Central government, central plus state to state government. So, and they should have added. A government company, if they are holding any shares in the central government holding shares in government company, if they are also investing, you should add that. Have they given that in the definition? No. Then why are you adding? Agreed? Pakka? Yes. Exam question, remember, Pakka people will go wrong there. Next one is called foreign company. What do you mean by foreign company? A company which is incorporated outside India but has a place of business in India and carries on some business activity in India. We call such company as a foreign company. Section 8 company means what? A company which is incorporated for charity, religious, science, arts, commerce, all these things. Two things that can come there. Always remember, a company, Section 8 company can never declare dividends and they cannot share profits. Agreed? And if at all you have done anything fraudulent, whatever is a license given to you to operate as a Section 8 company, that will be revoked. And what will happen to the existence of Section 8 company? Central government can tell that I can merge you with another Section 8 company, or I can wind you up, or I can convert your status from Section 8 company. Anyways, you are not doing charity. Convert yourself to a private company and do business in an ethical way. Why do it in the Section 8 company form? Correct? Okay. Next one, incorporation of a company. How to incorporate a company? We file one form, people. That's the main thing, called as SPICE plus. SPICE stands for Simplified Proforma of Incorporating Companies Electronically. What is this plus? So over a period of time, there was amendments that took place to the form. Changes. The changes was notified in the form of plus. We file all these forms with a person called as registrar. Correct? Now, depending upon the type of the company, we will always have, if it's a OPC, the name will have OPC Private Limited. If it's a public company, it will have the words limited. If it's a private company, it will have the words private limited. Correct? And accordingly, number of members are 1, 2, 7. We'll file an application. SPICE plus, that's application. You will give all the details there, shareholding details, directors details, MOA, AOA. You will file everything with them. If all the documents are fair, correct, proper, and people, that is when ROC will issue something called as Certificate of Incorporation. From that day, your company comes into existence. Agreed? Hello. What do you know a small company? Small company. XYZ Limited has a paid up capital of 3 crore. They have a turnover of 40 crore. Is this considered as a small company? Yes or no? Exact 40. Exact 40. So is it a small company or not? Now what is the definition of small company? A company. A company. A company. A company. Is it a small company? No. XYZ Limited is a public company. Can they be called as a small company? Ille. Correct? So people, a company other than public company having a paid up capital not exceeding 4 crore, having turnover not exceeding 40 crore. And certain companies can never be called as a small company. Who are they? First one, subsidiary company, holding companies can never be called as subsidiary, small companies. What do I mean by that? There is a company called as, let us imagine, XYZ Private Limited. There is a company called as ABC Private Limited. XYZ Private Limited holds 51% of shares in ABC Private Limited. ABC Private Limited paid up capital is 1 crore. The turnover is people 25 crore. Is ABC Private Limited a subsidiary Is it a small company? Is it a small company? Yes or no? Answer is no. Because small company definition clearly tells holding company, subsidiary company, Section 8 company, statutory company can never become a Section 8 company, can never become a small companies. So in total, remember, 5 companies are excluded. Sorry, 4 companies are excluded. Who are they? 5 only. A public company, holding company, subsidiary company, Section 8 company, statutory company. Who is a statutory company here? Anybody na? Yaro no? ICI. 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 It's a statutory corporation. It's a statutory company. Even if your turnover is less than 40 crore, capital less than 4 crore, you cannot be termed as. Clear up. Hello. Okay, incorporation automatically done. If you give incorrect details and incorporate a company people, then what will happen? Pass an order for regulation of management of company including changes in MOA. Meaning people, we have filed fraudulent details with ROC to register a company. If registrar gets to know, what will he do? He will say, you directors come down, I will replace the management. I will tell who the directors has to be. So I can replace the board. Next one, I can make changes in the MOA, OA. ROC has that right. Next one, I can make the liability of the shareholders unlimited. Director, removal of name from ROC. This is also called as easiest way, strike off. When you were registered, we wrote your name in the register of companies. In that, we will strike your name off. I can even pass an order for winding up. What is the difference between strike off and winding up? Winding up is a lengthy process. It includes liquidation. Assets has to be sold. Whereas in strike off, the company has not yet started the process. It is in the very early stage. Easy to cut down the business when compared to the winding up. Winding up includes dissolution, meaning liquidation. Assets has to be sold. Liabilities to be repaid. Only then I can wind up. Hello? Such an order as it may deem fit. Types of share, equity share and preference share. Correct? Types of share. There can be two types of share. One is ordinary share, one is DVR share. What do you mean by DVR share? Differential voting rights. What do you mean by differential voting rights? Generally what happens? Correct. When one share, see, when normal share people will have one share is equal to one vote in a meeting. One share is equal to probably 1 rupee as dividend. But if a company gives this in a different proportion, let us imagine one share is equal to, or say for example, 5 shares is equal to 1 vote. But 5 shares is equal to say 10 rupees as dividend. When compared to a normal share, if we are treating them a little differently, we call such equity shares as DVR shares. One company which had DVR shares no longer has is called as people Tata Motors. Tata Motors had normal share also, Tata Motor had DVR share also. This year only they have called off. They have discontinued the DVR shares. Now they do not have it anymore. They had it almost for a period of 15-18 years. Now they don't have it anymore, but they had it till this year. Such type of shares is called as what? DVR shares. Next one is called as preference share. What do you mean preference? Having a preference. Simple. There are 2 students. I prefer one student over the other. So remember, for a comparison to happen, there should always be equity shareholder. Only preference shareholder can never exist in a company. Preference means what? I am giving some priority. Sir, priority means in what are you giving priority? In 2 cases, when I am paying dividends, first I will pay to him and then to an equity shareholder. Next one, when a company is going for winding up, first I will pay to him. If I still have money, I will pay to equity shareholder. So between 2 siblings, there is discrimination. You discriminate preference shareholders. If you are making discrimination, so remember always, only preference shareholder can never exist. Clear up? Okay, company's documents. There are 2 types of documents. What are the 2 types of documents? Moe only. So, what are the clauses of MOA? What will be there in MOA? I'll tell you. Object for which? There will be clauses. No, what do you mean by the clauses? In the class, we would have seen Infosys MOA. Just search Infosys MOA. You guys will get. You can see the actual document. You can see all these clauses. Clauses are nothing but paragraphs, people. That's all. The first clause will be name clause. It signifies the name of company and type of company. Private limited, limited, OPC. Next one, registered office clause. What does it signify? It signifies state, meaning address. Only state. Third one, object clause. Purpose of the company. Meaning Arivu's object clause. Education. Liability clause. It says type of company. Liability, unlimited, limited, guarantee. Capital clause. What is the maximum capital of the company? That is only called as authorized capital. Association clause, also called as subscription clause. Nothing but who the initial shareholders are. Remember, FII, simply telling, from here to here can be altered. This can never be altered in the life of the company. Subscription clause, until the death of the company, will be the same. If you look at Tata Steel, when they registered, who were the first shareholders, their names only will be there. So subscription clause is simple. Who are the initial shareholders, their names will be there. That's all. If you look at Infosys, you can see 7 shareholders, including Narayan Murthy, Nandan Nilekani. You can see their names. Hello? Okay. Next one, articles of association. What is AOA? Internal rules of the company. It binds the company and its internal people, directors. So the rules set for the internal regulation is called as what, people? AOA. Okay. In the AOA, there is a concept of entrenchment. What do you mean by entrenchment? Huh? What do you mean by entrenchment? Making the rules stricter than the regular rules. For example, people, to clear your CA foundation exams, how much you should score? 200. Individually 40. Now, people, for mock exams, when you are writing, what is your class internal passing marks? If tests are conducted in the exam, here also 40 only. Yes, sir. Now let us imagine, people, I'll come and say the passing marks for law is 50 inside the class. Why? What is the intention? You clear this. You will definitely clear this. So I'm making the rules applicable to us stricter, so that you will pass the bigger exam. Hello? Agreed? Now can I make it 30? Now this concept is called as what, people? I can make it 50. Allowed? Yes, sir. This concept is called as what? Entrenchment. Can I make it 30? No. Why? This concept is called as what? Ultra wires. If Act says minimum is 40, I cannot make it 30. Hello? Pakana? How do I do entrenchment of articles? Which type of company? Public company? For both special resolution. Or for public company something and private company something. Public company special resolution. Private? Very good. Public company you have to pass special resolution. Private company, if you want to entrench your articles, meaning if you want to make it stricter, remember all the shareholders have to agree. You have to pass unanimous approval. Hello? Exam point of view, important. Remember and go. Possible examination question. Okay. Last one, sir, doctrines. Tell me now, what is doctrines, sir? So we know, what are all the doctrines we know? Doctrine of ultra wires, doctrine of constructive notice, Dr. Strange, indoor punishment. So, ultra wires means what? Beyond the powers of the Kamani. What do you mean by that? You are not supposed to do something which is not mentioned in MOA. Now, simple object clause. Agreed? Now, imagine, people, in Arivu's MOA, it is clearly written we can do education. Now, don't you think? I'll tell you one very easiest business opportunity. There is one space in ground floor. Open one kiosk, cafe, small cafe. Give ready to eat snacks and coffee and tea, nothing else. and give yes this chips and chocolates. Regular evening, 6 o'clock, CA inter class, 150 students strength. And this class here, there are 4 classrooms. Let us take together is 150. Up employees, there are around another 60 to 80 people. Just to open something. Thank me later. Full business. Yes, sir. Pramod started thinking, sir, nice idea. He should have come earlier. Yes or no? Actually, no. Actually, try. It's good business. Permission. You're considering, huh? We can. That's the, huh? Tell me how much you will give me. Accordingly, you will give, huh? Nominal illa. Sleeping partner, okay. Oh. Huh? But for me, 70. Why that much, da? Hey, that much all don't want, da. Even as if you only will go and do tea. You will do tea, ah. Pramod? I will do and reel and send it to your parents. CA ambition. CA ಮಾಡ್ಕೊಂಡ್ ಬಾರ ಅಂದ್ರೆ ಕಾಫಿ ಅಣ್ಣ you became. What? Okay. So, Pramod has all crazy ideas. I'll give you even better idea, na. 75,000 rupees investment. Pakka money, huh? 75 pakka money. What is that? Invest 75,000. You will get something called as vending machine. No rent, no hassle. Just to keep filling stock. Coke, Pepsi. That's whatever damages intestine and kidneys. Put it. Wow, that's it. You put all of these. Full money. No rent, nothing required. Correct, no? Huh? Nothing. I'm saying easiest way. Correct. Electricity, few expenses are there. But easy maintenance, no? Full money. Trust me. Sir, bitpudi, stay bitpudi. First tell us what else is there. We are more interested in that. Correct, no? Oh, yes. 100%. Always in for partnership.
Nominal partner.
Selfish, da. She will make so much money. For me, little also she is not giving. Then for me, what is enough, da?
Yeah, popularity, free advertising.
Give me money, nothing else. There is one saying, take money, everything follows. See, long time and all it was there, people. If anyone in your life, remember, anyone comes and tells you, I'm doing this only for passion, including teaching. Anyone, you might have met 500 teachers. Anyone tells you, we are doing teaching for passion, don't believe. Such things does not exist. Yeah? See, such things can never exist. Of course, teaching is a passion. I'll not deny it. But for a bike to run, petrol is important. I cannot say driving is passion. I know I can drive, but I need to go front also, no? I can't just sit in the same seat. Yes, same thing. Fuel is yum. Vitamin yum. Money. Money irka, yellamo irko. Money illaya, ennamo illa. Correct, huh? One great saying also, something like that also they say, no? To become a philosopher, for that also first you need to achieve it seems. First you achieve, then that is when you can become philosopher. If not, they will say mad. There's a difference between, see, the only difference between drunkard, mad and a philosopher is the status. Or else you tell me, a person whoever has drunk full, Paramatma, you go and meet with him. You speak to him for half an hour. You see the clarity in life he has. He knows what his life is for. He has full clarity. I'll drink, I'll go home, I'll sleep. He'll not cause any harm to anyone. Of course, he can't walk straight, but rest and all he can manage on his own. That much of clarity who will have? And you see the gems that comes out of his mouth. Hey, gems andre ido. I'm saying words. Movie, very movie. Huh? Huh? So much of clarity will have. Yes or no? So man, huh? Let us do something. Allah Guru. Correct, no? We'll do something.
Yes, sir.
What?
See.
CA foundation, no? Matte do foundation first. Huh? Okay. It means beyond the power of company. Impact. Such contracts shall be void. Hence, neither the company can be sued nor the company can sue the third party. So, what do you mean by that? Now, say for example, whatever I told you, in our object clause, we say we can do education. But our object clause, now what I'll do, there is a wonderful opportunity to start one cafe, tea, and we can do one fried rice. Generally, if you mix it, 50 rupees. If it touches roofs and comes down, 100 rupees. Correct? No, takak. And you have to keep making sound. Taka, taka, 150 rupees. Now, people, now what I'll do, I'll start a cafe. The first question we will ask you is, what does your MOA say? Education. Now, any contract I enter for cafe, I might have purchased raw materials, I might have entered into a rental agreement with my owner. All these agreements are considered as a void. It will not bind the company. Then whom will it bind? Whoever entered into the contract, they will be personally liable, not the company. Sir, let us imagine, what does ArivuPro's object clause say? We are into education. Now let us imagine, sir, one creditor gave money to ArivuPro. For what? Let us imagine, we borrowed money for the cafe business. He believed in us and he gave money. But we used that money for some other purpose. We had some other debt. We used this money to repay that debt. I used this money to repay one more debt. Now when this person is asking back money, we are saying ultra wires da. We cannot borrow money for cafe business. Why did you give? We will not repay. Now you tell me, will this bind the company? Should we repay the debt? Should we repay? Yes or no? You will have to repay. Remember, if at all the company has made use of that money, you have used that money to repay one more debt. Correct? Ultra wires is correct. It does not bind the company. Then why did you use that money? Using that you repaid one more legal debt, right? But if you had used that money towards your cafe business, now that people, you were not authorized. That in that case, the directors, whoever took that loan, they will be personally liable. But if company has made a benefit out of it, you have used that money, you will be liable to repay. Even though it is a void agreement, you made a benefit of it. Hello?
Yes,
Agreed? Now this is only called as what people ultra wires transactions, void ab initio. Clear? The next type of contract is called as what people doctrine of constructive notice. What do you mean by doctrine of constructive notice? Whatever documents I'm talking about, people, all these documents sit in the public domain. It sits on MCA website. Anyone wants, they can download, they can see whatever is there. It's not a rocket science. Agreed? Yes. Now people, anyone who is entering into a contract with the company, it is assumed that you have read all the documents in the public domain, whether you know it or not. Remember people, ignorance of law is not an excuse. Me driving in Vietnam, Anna please, bitpidi. Did they leave me? No. Ignorance of law is not an excuse. You will be liable. Agreed? So when a person is entering into a contract with the company, he cannot say, now the creditor in the previous case cannot say, sir, I did not know that their MOA says cafe business. I gave it in a very good faith. we will say whether you read it or not. If you are giving money to the company, if you are entering into an agreement with the company, you are assumed to have the knowledge of MOA, AOA. You are assumed. Hello? Understood all of you? Okay. Next ones are indoor management. What do you mean by indoor management? Huh? Hello? Whatever happens within these 4 doors. Now one lady walked. I'll call her and I ask how to do cafe business. She will tell, but we discussed, no. Then can't she tell that? She was not in the company. Macha, just like that, in general meeting, we will not allow the outsiders. Not every information is there in the public domain. If at all the information is available in the public domain and you have not read it, then constructive notice will come. Sir, what if the information itself is not there in the public domain? Then people, we call it as indoor management. Remember, doctrine of constructive notice protects the company from the outsiders. Sorry, outsiders from the company. Doctrine of indoor management protects the outsiders from the company. Hello? Pakkana? Allah, yes or no, something. Last ones are exceptions to doctrine of indoor management. First one is the case law. Actual or constructive knowledge of irregularity. Simple people. Doctrine of indoor management will not apply if you knew about that irregularity. What do you mean by that? Okay. These things we'll do up directly in the case only. We'll cover in the case law part only. Because I have to anyways explain the cases. If not, that entire concept only I can't explain. That part, it is linked with case laws. We'll see with case laws only. Hello? Okay. That's your company's act. Hello? Okay. Next we'll do of negotiable instrument. If you guys want, take a quick 5 or 10 minutes break and taka come back. We'll finish off negotiable instruments and LLP. Maximum another maximum 1 hour. A break, if you want, go back, go for 10 minutes and come fast. But in between, let us not break it. Go. Yes, people, next one, easy chapter. Let us do it of LLP. Very easy. I told you already the weightage. Very important from exam point of view. Read and go. Don't leave it. Yes, sir? Okay. Now, what do you mean by LLP, people? LLP stands for Limited Liability Partnership. Now, why should someone choose LLP? That is the reason. Reason is, people, they enjoy the characteristics of partnership also. They enjoy the characteristics of company also. That's why we call this as a hybrid instrument. It's a hybrid of company and partnership. Whatever are the characteristics you saw in a company, all that is there in LLP as well. What are the characteristics we saw? We saw separate legal entity, limited liability, perpetual succession, artificial person, and common seal, which is again optional. And what else? Now, for example, the number of members in public company. What are the number of members in public company? Minimum is 7. Maximum is unlimited. Remember, in LLP also, the maximum number of partners is unlimited. You can have any number of partners. There is no limit at all. Now, what other characteristics are there? Now, in a company, we used to file all the documents with registrar. Cut, copy, paste. Everything will apply. Sir, company was taken care by ROC. Who takes care of LLP? Same person only. Registrar of companies only take care of that also. Cut, copy, paste. Whatever is there in company, everything applies to LLP as well. Now, why should someone choose company in LLP? Company, people, is more strict. It does not have flexibility. If you want maximum flexibility, you should always go with partnership. Maximum flexibility, because no governing, even registration is also optional. You need not have to file anything. No one comes and cares what is happening. So literally everything is optional. You need not have to file any forms. People will not even know whether you exist or don't exist. That's the best example. Full on flexibility, partnership. But there is a risk. What is that? Anything happens, liability is unlimited. You will lose everything that you have earned. Now, in case of Byju's or in case of Videocon, all this, what is helping the founders? The shield. That is only limited liability. Agreed. Sir, but I want some characteristics that partnership also has. What is that? Flexibility. Here everything you have to follow Companies Act. But in LLP deed people, in LLP, just like partnership, you will have LLP deed. Whatever your LLP deed says, you can follow that. Flexible. Sir, in partnership, there are partners. Here also there are partners. In company, that power is split. No. If you actually look at the difference between company, LLP and partnership, in company and LLP, the nature and characteristics are almost same. Correct? Huh? Sir, here, who are the owners of the company? Very good. Correct. Shareholders. Who are the management of the company? Who takes care of management? Board of directors. In the case of partnership, everything is partners only. In the case of LLP, who are the owners? Partners. Who are the management? Who take care of management? Remember, partners only. There is nothing called designated partners who take care of management. Designated partners just to take care of compliances, GST filings, legal filings, IT returns. Only that part they are responsible. Running the company, running the management is with all the partners. Hello?
Yes, sir.
Okay. Now, sir, what else is the difference? What is the maximum number of shareholders? We saw here. Maximum partners we saw here. Here it is unlimited. Sir, remember, can there be a foreign company? Answer is yes. Can there be a foreign partnership?
No.
Answer is no. A foreigner cannot invest in a partnership firm. But can a foreigner invest in LLP? Answer is yes. Same like company, foreign company is there. There is foreign LLP also. A LLP registered outside India, which has a place of business in India. We call that as foreign LLP. Sir, here we call it as capital. Here we call it as, meaning here we call it as share capital. What do we call it here as? Contribution. Understood? Huh? Yes, sir. How many minimum partners should LLP have? Minimum is 2. Now there is one more type of partner is called as, what is he? Designated partner. How many minimum designated partners the LLP should have? So minimum people required to start LLP, how much? How much? Minimum people to start, how many people required? The 2 partners only will become the 2 designated partners. Agreed? And remember, in these 2 designated partners also, one should always be resident in India during the financial year. OPC is previous financial year. LLP is during the financial year. So out of 2 designated partners, at least one should be residing in India. Why? Accountability. We should catch hold of someone at any given point of time. Agreed? No. If something happens, everyone runs away. Then whom shall we file a case on? We will all get it done by this person. So designated partner, one person resident in India is mandatory. Agreed? Hello? Sir, when will this person be called as a resident? You should stay in India for 120 days during the financial year. Meaning in the current year you should stay. It's an ongoing basis. Next year also same thing. Next year also same thing. As long as the LLP continues, you need to satisfy this condition. Hello? Agreed? Okay. So what are the characteristics of LLP, partners, difference? Okay. Yes, sir. Features, sir. Is LLP a body corporate? What is the definition of body corporate? What and all is considered as body corporate? Company, foreign company, remember, all these people together are called as body corporate. They can ask you a question, remember and go. Hello? Okay. LLP is a body corporate. It has perpetual succession, separate legal entity. I told you, same characteristics as a company. It has a mutual agency. Remember, there are 3 partners. If one partner is going and signing any contract, just like partnership, in partnership, what is happening? One partner goes and signs. He is binding all the other partners. No. In LLP, that is not the case. He can never bind the partners personally. You can only bind the LLP. For whatever contracts you enter, LLP is liable, but not the partners personally. That's the difference. So mutual agency is there. Any partner can represent the LLP, but he cannot represent another partner. So whatever one partner does, the other partners are always safe. They have no risk. Hello? Next one, LLP agreement. Just like partnership deed, here it is LLP deed. It is considered as artificial legal person. Common seal, mandatory, yeah? Same thing. May. Limited liability, yeah? Minimum members how many? Maximum unlimited. Compromise arrangement not required. Leave it. Conversion into LLP. Can a private company convert into LLP? Possible. Can a public company convert? Yes, anyone can convert a unlisted public company, private company, OPC, partnership firm. Anyone can convert from one form to LLP. If you think LLP is beneficial to you, come and convert. It is okay. We will allow you. We don't have any problem. Hello? Which one? Meaning you cannot do a Section 8 activity under LLP. That is not possible. That is not possible. In Section 8 company, there can be one question. What is that? Can a partnership firm be a shareholder in a company? Can a partnership firm be a shareholder in a company? Not possible. Only exception is in Section 8 company, partnership firm can be a shareholder. Remember this. They can ask you somewhere. Correct? Yes, sir.
If a company can be a shareholder in another company, then why not a partnership?
Partnership firm is not a separate legal person. No, they do not exist.
In case of LLP,
LLP can be a shareholder. LLP is a body corporate. LLP can be a shareholder in one company. That is possible. Yes, agreed. Yes, sir. A partnership firm, not LLP. Partnership firm cannot be a shareholder in another company. I cannot hold shares because legally I don't exist. I'm not a body corporate. So I don't have existence of my own. But Companies Act has specifically given an exception. That exception is a Section 8 company, a partnership firm can be a shareholder. So in the name of partnership firm, you can invest money in Section 8 company. We allow that. And nowhere else we allow. Dividend will not be paid. That's why the whole purpose is that only, no? It is not for money. That's why we are allowing. Agreed, huh? Hello? Next one, business for. Same thing. Management of business. Who is managing the business? Remember, never write designated partners. Investigation, just like a company, central government can conduct investigation on LLPs. E-filing of documents, I told you. There we filed every document. Here also you have to file, mandatory. Foreign LLP concept exists here as well. LLP registered outside India has a place of business in India. Incorporation of LLP. How do we incorporate LLP? Same way. However, you guys did the company. The minimum 2 partners along with the names of designated partners, you have to file a form. The form is called as people. Form Philip. Form of incorporating limited liability partnership. You file it with whom? You file it with registrar only. If registrar is satisfied with whatever information you guys have given, registrar will give you certificate of incorporation. One form is important here, that is only called as there shall be a statement filed. They can ask you this question, remember and go. So along with the Philip form, I have to give one statement, it seems. What is a statement? Meaning a declaration. Whatever we have filed, all the documents, information we have filed is true. There shall be filed along with the incorporation document, a statement. It may be either who should sign it. An advocate can sign it, a CS can sign it, CA can sign it, CMA can sign it, who is engaged in the formation of LLP. So we should sign. And by anyone who subscribed his name to the incorporation document, that means what? A partner. So technically people, let us imagine one CA has to sign and one partner has to sign. That whatever is the requirements under the law, we have followed everything. Dear registrar, we are giving like a personal guarantee. You guys can think, why are we coming here? Then why are we passing these exams? Just out, exactly. But remember, this passion comes with a little expense. If you do some mistake in job, maximum they'll remove you. Here, direct jail. Imprisonment is the penalty. Why? I'll tell you that also. I'll tell you. Imagine something like Kingfisher, that scam happened. I don't know if you guys know. The reason for Satyam scam, I think you would have heard of. Why did Satyam scam happen? Internal auditors did not do their job properly. Yes, that means what? Every year you have been filing financials with wrong details. Who should have checked it? That is also there. That is what I'm saying. Now you can just say, right, sir, bad time, sir. It's okay. I'll resign and go. $2 million penalty, suspension for 3 years. It can even result into debarment of your certificate. You can be imprisonment up to 10 years. You'll see Companies Act. There is one entire chapter on you. Yes, sir. Then that's how it is. Why did we do it? Agreed, Macha, remember, why is your sign there? Government only one person. For Karnataka, only one registrar is there. Like that, every state has only one registrar. There are some exceptions. We don't want it. So one person, can he check all the details? No. That is how our profession took birth. We promised, our institutes, our 3 sister institutes promised government, you don't worry, we will reduce your burden. We will check and file. You just take it blindly. Now, Macha, when he is taking blindly, if something goes wrong, they will make us blind. 100%. And remember, people, a criminal record on us is an life end. Correct, no? You remember so many forms you will be filling. In every place they will be there. Were you arrested for any reason? You will have to put a tick mark there. In which job will that? See, did I tell you did a mistake? Did I tell you did a fraud? It might be negligence also. You are liable. Come back. Okay, registered office of LLP and change therein. Every LLP shall have a registered office. If you change the registered office also, you are expected to communicate the change. Agreed? After the LLP is registered, you will have a right to sue, be sued. You can acquire, you can hold property in your name, company, common seal. All that is cut, copy, paste. Yes. And one thing that is important is change of name. Agreed? Remember, LLP has a name XYZ LLP. Can the LLP change its name any given point of time? Same provision applies to even company also. I am telling the same provisions both together. You both can change, company and LLP. They can change their name in two ways. One is voluntary. Whenever they want, they can change. Example, there was a company called as Zomato. They changed their company's name into. Don't tell me, don't know. 1 year I thought. Said no, sir. In my mobile, it is still showing Zomato only. That's their trademark. The name of the company has changed. Yes, sir. So their name is Eternal now. Eternal, Eternal. Eternal Limited. That's the name of the company. I get in the point. So they can change. It's a voluntary name change. Whenever they want, they can change. So the next one is called as what? Mandatory. Someone tells you to change. You have to change. You don't have a choice. Sir, when will this happen? Correct. When there are two LLPs or companies or registered trademarks with similar name, they will come and say, sir, that second company is same as our name. Can you please tell them to change? We will go and complain it to the central government. Central government, if it is convinced, what will central government do? Central government will pass an order. AU LLP or AU company. Your name is similar to that person's name. Why did you register with this name? Change first. You will be given some time to change. How much? You will be given 3 months time to change from the date of the order passed by central government. If you do not change within 3 months, people, central government only will allot you the new name. And the new name will not be nice. You guys will not like it. The name will be Central Government's Order Not Complied. Serial number 2025 Limited. That will be the name. And remember, new certificate of incorporation will be issued. So you will get that. The moment you get a certificate of incorporation, you are liable to change all your documents, including the name board in front of your office. It's a legal requirement. You have to put it. See how it will look. Correct? No. So to avoid that, they are telling you, better you only change it. Sir, after they giving a name, can we further change it? That is possible. I'm not telling you cannot change. But at least one day you will have that name. Yes, sir. Sir, who can go and complain? This company one came and complained. No, that company's name is similar to me. That LLP's name is similar to me. This person should go to the court within 3 years from the date of this company two's incorporation. So the dummy company gets incorporated. No, within 2 years I need to go and complain. Within 3 years. If I do not go within 3 years, I lose my right to go and complain forever. Hello. When you get time, search on MC. I don't know if you guys have all done that MCA search and all. No? Okay, leave it. Done. That's your LLP. Any doubts? Hello. Okay, done. The last part, sir, let us come to negotiable instruments. Now, people, what is negotiable instruments? Negotiable instruments, correct? What do you mean by negotiable instruments? The word negotiable means what, people? Transferable. An instrument which can be transferred, people, any number of times until the date of maturity is called as what, people? A negotiable instrument. So, for example, A borrows a loan from B as a security. B will demand, hey, give me some document that so that if you do not repay me the money, I should have something to file a case on you. A will write one letter and give it to B. Macha, thank you for giving so much of money. Anana, I need to pay you 5 lakh at the rate of Anana, I will repay it to you after 6 months. Thanking you, yours lovingly. Will write that letter. Now, people, this is only called as what, people? Promissory note. Agreed? Of course, it will not be like that, but yes, more or less. Clear? Hello? Okay. So, sir, what are the characteristics of negotiable instrument? What are characteristics of negotiable instrument? It must be in writing. It should be cash only. It cannot be any other thing. It should be money only. Nothing else can exist. And it should be signed. It should be transferable. It should be transferred. I cannot write this letter and I can only not keep it. I have to give it. Agreed? It should be free from defects. Okay. Now see sir, essential characteristics sir. It should be in writing, signed, it should be freely transferable, it should be unconditional. I cannot say if Salman Khan gets married is when I'll give you the money. Yes sir. So can it not be conditional? Can it be conditional? It cannot be conditional. Remember, conditional is possible if it is certain. Meaning, say for example, this is uncertain or certain? Okay, we'll let it, I don't know. So, if it is certain, you can have it. Certain is what? I will pay you the money by the sunrise or the sunset. It's a conditional event, but it is certain. You know that sunrise will happen, hopefully. Yes, no. So, that is conditional, it is allowed, it is agreed. Next one is cause. It has to be to pay money only. Instrument must be delivered. Remember, I enter into a promissory note. I'll give you 5,000 tengin kai, coconut. This cannot be a promissory note. It has to be cash. If cash is not involved, it cannot be called as negotiable instrument at all. First of all, what is the definition of negotiable instrument? Definition of negotiable instrument. Very good. There is no definition at all. And that also you guys will define. That's why I like students. Understood? You will have answer to anything. Anything and everything. Negotiable instrument is not defined at all. It only says what are the different types of negotiable instruments. 3 irko. One is promissory note. One is bill of exchange. Check. Okay. Now what do you mean by promissory note? What are the parties to promissory note? There are 2 people. Who are they? Maker. Second one is called payee. Who is the maker? Technically the debtor. The person who promises to pay the money is called as maker. Payee means what? The person to whom we have made the promise is called as payee. Correct. Characteristics will be similar to whatever is of negotiable instrument. It should be in writing, it should be signed, it should be transferred, it should be unconditional, it should be definite, certain, cash only. That is all same. Katta, copy, paste. And remember one thing, all these instruments has to be mandatorily stamped. Yen sir, put it on the ground and just stamp it. How many times you want to stamp it, sir? Tell us, we will do. Stamp means what? Stamp means what? Means putting stamps. 2 rupee na? 1 rupee paper. Huh? There 1 rupee paper, sir. What is it? 1 rupee paper? Yo, Pramod, I like the way you are playing this dumb charades vocally. Okay. Now understood, Stamp means what? Revenue stamps, it's called. Postal stamps. That only, no? That is Gandhi Jatan will be there, no? Note Allah. That only, sir. Yes, So it can be that. That is called as revenue or postal stamps. Different types of stamps exist. Today we enter into e-stamps. We don't have postal stamps today. We don't follow it. We follow e-stamps today. Hello, understood? What do you mean by promissory note? It is an unconditional undertaking. Undertaking means what? Promise. I am making a pinky promise. I am saying, sir, I will pakka pay the money. Promise on you. That's why it's called promissory note. No, undertaking means what? Someone is taking an oath. I'll pakka pay, sir. Guarantee. That is only called as what? Promissory note. It is an unconditional undertaking signed by the maker to pay a certain sum of money. Certain, see. It cannot be vague. Only to or to the order of certain person or bearer of the instrument. Let us see if it is there here. I hope you guys have seen promissory notes. Yes, sir. Yesterday only I wrote one. See, promise note. Pramod. அதுதானா? Finally. People, this promissory note was made in 16th December 1926. Okay, 20,000 rupees it seems. We can buy half of Bangalore that time. On demand, we promised to pay at Imperial Bank of India, Rangoon, to OAOKCJ Karuppan Chettiar Anna, or order for value received the sum of rupees 20,000 only with interest from this day at the rate of 6.5% per annum, and this person has signed who? PN LV Somasundaram Chettiar. You don't know how to read Tamil? Then read English. You thought I had special talent, huh? எப்படியே? Yes, Somasundaram Chettiar. Now this person has signed this promise note that I will pay to whom? OAOKCJ Karuppan Chettiar. By his attorney. That means someone has acted on behalf of me. Whose liability it is principal? Technically it is nothing but principal agent relationship. See, in one document how many relationships are there? Correct? Hello? Got a fair idea na? No, it has to be mandatorily stamped. This is the meaning of stamp. Clear? Hello? Off late, I mean that time people, you used to get these as a predefined documents in banks. Banks used to give this. If you see it only the dash has been filled. That were the days. We used to get a ready-made thing in banks. We used to just take it. If you see, there will be registration numbers also over it. So those times it used to exist. See, if you see, Imperial Bank has signed it. It's a seal. So it's a bank official promissory note. If you see, everything is happening inside the bank. That's why the place of payment is where, see, to pay at Imperial Bank of Rangoon. Place of payment. Hello? Got a fair idea? Yes, this is the meaning of promissory note. Okay, the next one is called as what people? Bill of exchange. What do you mean by bill of exchange now? It is an unconditional order. How does a bill of exchange come into picture? There will be a party. There will be a party. A person purchases something on credit. So imagine I supply raw material and I give him credit period to repay. But what is the guarantee that he will repay? So to be safe, what will I do? I will tell him, people, do one thing. I will draw one instrument and give you. You sign it and send it back to me. So people, I will only prepare the bill. I will give it to him to sign and send it back. The bill which is prepared by the creditor only or the seller only and given to the debtor to sign, to see and send it back is called as, people, bill of exchange. Clear? Yes, sir. In bill of exchange, how many parties exist? It can be 3. One is called as drawer, drawee, payee. Remember, drawer and payee can be the same person, or drawer can tell someone else, pay it to him, don't pay it to me. That is also possible. The person who draws the bill is called as drawer. The person who needs to make the payment is called as drawee. The person to whom the money is given, entitled, is called as payee. Agreed? Okay. Parties, drawer, drawee, payee. Acceptor for all, this is not there for us, leave it. Holder. Okay, come to classification of negotiable instruments. What do you mean by classification of negotiable instruments? There are different types of negotiable instruments means. What do you mean by that? Negotiable instruments can be classified based on parties. First one, if at all the party's name is not mentioned on the instrument, what type of instrument we call it as? Bearer instrument. Sir, the name of the parties are clearly mentioned. We call such instruments as order instrument. OA, OK, CJ, Karuppan, Chettiar, Ano. Now what is this called as? Order instrument. When the name is clearly written. Agreed? When that blank is not filled, it becomes a bearer instrument. Based on validity, the instrument can be classified into two things. One is called as inchoate, one is called as ambiguous. What do you mean by inchoate? Inchoate means, people, it is not complete. The person delivers a blank instrument to complete with appropriate amount up to the stamp value of the instrument. Now what do I mean by that? Now let us imagine, people, there is a person, okay, there is Mr. A. Mr. A's, say for example, daughter wants to join ArivuPro for classes. For how many classes, we are not sure. She wants to try first one subject. So for one subject, let us imagine, people, the fees is, I don't know, how much da? Okay, 5,000 rupees is the fees for one subject, let us imagine. Now people, the father has to make the admission, he needs to make the payment and go. They are from a different place. Now how much payment should be made? Now people, if it is one subject, it is 5,000, 4 subjects, 20,000. But as on today, the daughter is unsure. She wants to try. If it is okay, I will continue all 4. If it is only one, I will see this. If it is not working, I will go back. Now people, what will the father do? The father will say, well, let us do one thing. I'll do one thing, I'll sign one instrument and I'll give along with the stamp papers. Because stamp paper is mandatory. It will always be a percentage of the total amount. Now for example, if you see that for 20,000 rupees, they have given 4 Anna. Let us imagine 4 rupees. To keep it simple, let us do one thing. For 20,000 rupees transaction, let us imagine 100 rupees is a stamp paper. We have to take stamp duty. We have to pay to the government and we need to get the stamps. So what I will do, Mr. A will take a promissory note. He will clearly write to ArivuPro and I will leave the amount blank. I will not fill it because I don't know whether it is 5,000 or 20,000. So I will leave it blank. And what I will do, I will affix stamp. How much? What is the maximum possible? 5 into 4 subjects. So the maximum amount possible I need to pay is 20,000. So father will pay stamp duty for 100 rupees and he will affix it here. Clear? Now this is given to ArivuPro. Hello? So is the instrument having the amount? Now people, I came and I taught you for the entire year. I've taught. I'm done. Now my salary is how much? 20,000 rupees. Now what will I do? I'll come and say my assignment is over for the year. ArivuPro, please give me my salary. Now what will ArivuPro do? Sir, do one thing. We have this instrument. You only take this. You go and encash it with the father. So they will endorse the instrument in my name. They will turn the page. They will write pay to Mr. Sai. They will sign it and they'll give it to me. Now what did this daughter do? The daughter joined only one subject and she did not continue. Now people, you tell me, how much should the father pay to ArivuPro? 5,000. Now what is my salary? Now I went and I gave this promissory note to the father. Sir, please 20,000, can you please give it to me? The daughter was there only. She said, Papa, no 25 only, don't give him 20. Now people, you tell me, how much can I recover? 20 or 5? I almost explained you Bahubali story. Hey, Abba. 20 5,000 25,000 yaar. 20? Now people, from father I can take only 5,000. Remember people, who is this person? This person is called as people Holder in due course. Kaun hai holder in due course? Holder in due course is people. My God. Holder in due course is like in this chapter, God ano. We will never disrespect God. Now people, holder in due course is like that. Meaning what? Who cares what has happened? On the document, what is the stamp duty? 100 rupees. 100 rupees is for how much money? For 20,000 it is 100 rupees. No. The father will have to pay the entire 20,000 rupees to me. Why? Because I am a holder in due course. What do you mean holder in due course? A person who gets an instrument written in his name before the maturity in good faith. Do I know all of this? I don't know any of this. And I earned this instrument. I did not get it free of cost. ArivuPro did not gift it to me. I earned it. In this case, what they are telling you? The right I get is called as people, holder in due course. I can recover the money up to the value of stamp duty. Hello? Option number first scenario, understood? Second scenario, sir. I went ArivuPro. They said, sir, very good job. We are congratulating you. We are giving you a gift. What is a gift? They gave me that promissory note. Why are they giving it to me, people, as a gift? Now I took this to Mr. A, father. I'm asking for money. Now you tell me, what is the maximum money the father will pay me? The maximum money now. I'm not a holder in due course. I did not get the instrument for value. I did not earn it. I got it free. Now people, the maximum liability of the person, that is Mr. A, cannot be more than what he has legally supposed to pay. How much he is legally supposed to pay? 5,000. That's the difference between holder in due course and a normal person. You earn it. You always have a better right. You get it as a gift or a free. You do not get that right. This is the concept of holder in due course. This is the concept of inchoate instrument. Understood? Hello? Pakka? Done. Next one is called as ambiguous instrument. What do you mean by ambiguous instrument? Whenever there is a confusion between whether it is a promissory note or bill of exchange, we call such instruments as people ambiguous instrument. You can consider it as either a promissory note or a bill of exchange. We consider it as a ambiguous instrument. At the option of the holder, whoever has the instrument, he will have a choice. If you want, you consider it as promissory note. If you want, you consider it as bill of exchange. When will it become like that? Always remember, a self-drawn bill. In bill of exchange, what happened? A drew the bill, he gave it to B to accept and give it back. It is drawn on someone else. But instead of that, if A draws the bill on himself, they are called as self-drawn bills. I am telling, I will pay Mr. B for so and so amount. Now what happened? It is looking similar to a promissory note. When there is a self-drawn bill, it will resemble a promissory note. That is when it will be called as an ambiguous instrument. When I draw a bill on myself, so when there are only two parties now. So ambiguous instrument is nothing but an instrument which has a color of promissory note also, bill of exchange also. The holder has a choice to choose. However he wants, he can choose. Once you choose it in one way, all the rules of that instrument will apply. Simple? Hello? Next one. Based on place, the instrument can be classified into inland or foreign. Important from exam point of view. What do you mean by inland instruments? Inland instruments means what, people? Remember three conditions. First thing, it should be drawn in India. Sir, the first condition only not satisfied. Directly it's a foreign instrument. Hello? Okay. Sir, it is drawn in India. But sir, where is it payable? Is it payable in India or Australia? If it is in India, in these two conditions, any one is at least satisfied, then it is an Indian instrument. Sir, what do I mean by that, sir? Let us imagine, it is drawn in Chennai. but it is payable in Singapore. Who should pay? The person residing in Singapore, he will pay. First condition satisfied in India. Bottom both conditions not satisfied. You will call this as foreign instrument. Hello? Let us imagine drawn in Chennai, payable in Singapore, but where does the drawee? Who makes the payment? The person who makes the payment, he resides in Bangalore. Inland instrument. Sir, the bill is drawn in Canada. The bill is drawn in Canada. Don't check anything else. If the bill itself is drawn outside India, then no matter what, it is a foreign instrument only. Hello? That's all. This is inland instrument. This is foreign instrument. Clear? Okay. Note. The foreign instrument is regulated by the law of place where he made the instrument. If bill is endorsed, the law of place where the instrument is made payable. What do I mean by that? Let us imagine A, B, C. A made the bill of, say for example, a negotiable instrument in Singapore. Sir, B is the person who has to make the payment. Let us imagine this person is the drawer. This person is the drawee. Now, where does the drawee reside? Let us imagine drawee resides in some place. Let us imagine Canada. Sir, if bill is endorsed, the law of place where the instrument is made payable. Now, what do I mean by that? Now, C, where does C reside? Let us imagine C resides in some place, India. Hello? Now, where was the bill drawn? Singapore. So, we know for a fact it is a foreign instrument. Now, what rules will apply? Singapore laws will apply, Canada laws will apply, India laws will apply, which law will apply? By default, wherever the bill is drawn, that rules will apply. So, Singapore rules will apply. Hello? Now, who should make the payment? B should make the payment. So, what I will do? I will take the bill to B and go. Or let us imagine, I will take the bill to B and go. Now, let us imagine, sir, if B dishonors the bill, meaning if B does not make the payment. Okay, let us imagine like this, people. A has transferred the bill to C. A has transferred the bill to C. The bill is endorsed now. They have transferred it. Now the rules will change. What they will say, if the bill is endorsed, A has given the bill to C. The law of place where the instrument is made payable. Now where will the instrument be payable? C will take the bill. C resides in India. If C needs to get the money, where should he go? I will go to Canada. Where is the bill payable? Canada. Now remember, people, once the bill is endorsed, the law of the land, wherever the instrument is made payable, that will apply. Now where is the instrument made payable? Canada. That is where the law will apply. Now Canada law will apply. Hello? 100%? So first, wherever the instrument is made, that is the law which will apply. If the bill is endorsed, they are telling you wherever the bill is made payable, that law will apply. Hello? Pakana. If B does not make the payment, now what will C do? Go to A. Pakka. Now which law will apply? If B does not make the payment. If B does not make the payment, which law will apply? C will take the bill and go to A node for making the payment. So where is the bill payable now? So which law will apply? Remember, exam, they may ask you this question. By default, wherever the bill is drawn, if the bill is endorsed, then wherever the bill is payable, that is the rule which will apply. Hello? Done. Drawn in a foreign instrument. Okay, based on time, there are two types of instrument. One is called as demand instrument, one is called as time instrument. Demand instrument means what? Demand instrument means what? Whenever the instrument is given, the instrument has to be paid. That is what? Demand instrument we call it, right? If you see, this example was also The first two letters only says what? Whenever you ask, we will pay. Or they will say, we will pay after 2 years. That becomes time instrument. Demand instrument means, if at all I come and give you the bill, you have to make the payment. That is called demand instrument. Sir, if I clearly write, the bill will be payable in 1930, that's all. It is called as time instrument. I have to wait till 1930. This time, even if I go and give it after 1 month, I'll get the payment. Hello? Then, okay. Sir, negotiation of negotiable instrument. How will you negotiate an instrument? Negotiate means what? Transfer. How will you transfer an instrument? Depends upon what type of instrument it is. If it is a bearer instrument or if it is an order instrument. Bearer means name is not there. When name is not there, you need not have to sign. Just to transfer it into their hand. Done. Because no one's name is there. Now, whereas if our OA, OK, CJ, Karupan, Chettiar, Anna, if he has to transfer, he has to turn the bill. He has to write, pay to Mr. Pramod Anna. And OA, OK, CJ, Karupan, Chettiar, Anna has to sign. Correct, huh? Yes or no? And I will sign and I will only keep it, huh? Illa. Remember, order instrument, sign plus delivery. Bearer instrument, only delivery. Agreed, huh? Hello. Yes or no, da? Okay, the last one is called as check. What do you check, da? The bill of exchange drawn specified bank, non-express drawn, includes estimate chunk. Okay, now what do you mean by this, da? People, check means what, da? Check means check. In check, people, check is also bill of exchange only, no? Check will always have 3 parties. Count. A, B, very good. C. Who is A? A is people, a drawer. Who is a drawer? The person who tears the checkbook. Rich guy. Who tears the checkbook. In that he will write, pay to this person who? C. Pay to him 1 lakh rupees. He is tearing a check and he is signing and giving it. The person who gives it is always called as drawer. Drawer. The person who tears the checkbook and gives is called as a drawer. To whomever the money is entitled, whoever gets the money is called as payee. Always remember, in the bank, who will make the payment? Always the bank makes the payment. So the drawee in a check is always a bank. Hello? And check is also a bill of instrument. It's a bill of exchange only. Of late, physical checks are also fading away. They are coming up with electronic checks, meaning some things which can be authorized by digital signatures, OTPs, etc. That's where they have included checks in electronic form. Yes, sir. And next type of check is called as truncated check. Truncated check is nothing but people a scanned check or a Xerox copy. In our easy language, I am telling you. Why will people take Xerox of a check? For movement. Now you are giving the money to one bank. C is going and depositing the money in ICICI Bank. But where is A having an account? Let us imagine Axis Bank. Now one bank will go and collect the money from another bank and come and deposit it. So the checker internally will have lot of movement. What if the check gets destroyed? You know how we treat documents. How do we treat? Parota. Correct, no? I love you, Janu. There only we will write. I have got notes with Gandhi Tata being full sketch and all they have done. What if the check happens the same thing? Gets destroyed. That's why what they do. They transfer it, they scan it. The scanned copy is only called as what? Truncated check. Understood? Types of check. One is open, one is closed. Alva. Cross the check. Open check means what? I go and give the check in the bank. The check will give me the money there only. They will give me physical cash if it's an open check. Cross the check means what? It's an instruction to the banker. Anna, don't give cash, sir. Only do bank transfer. I have given you the account number in the checker. Deposit the money to that account. Don't make the payment in cash. So much I can tell to the banker. Yes, how? By marking 2 lines. If 2 lines are marked on the checker, it's an instruction given by the drawer to the banker. Don't make a physical cash payment. Transfer the money to his account. So now, even if you lose it, it's okay. Whoever gets it, the money will be transferred to that account only. That's why crossed checks are always safe. Hello. Parties done. Last one, sir, check. Whenever there's a check bounce, how do we handle this case? If there's a check bounce, first drawer gave the check to payee. Why did we give a gift or earning? Remember, gift, the section is dead end. Check bounce case can never come in the case of gift. Inheritance, it can never come. You will get a right to fight check bounce case only if it is an earning. That's what it's called as legally enforceable debt. What is the returns here? Gift to donation and security is not covered under the section. Correct? Hello. Yes, sir. Okay. Tore it, gave it to the drawee. To the payee. Anamon will, what will he do? He will come, he will present the bill in the check in the bank. Of course, I have to present it within the time before it becomes stale. The validity of the check is 3 months from the date mentioned on it. If I don't give it, it becomes a stale check. So within that time, I have to mention, I have to go and present it. If at all money is there, they would have made the payment. Of course, money is not there. That's why what is the bank doing? The bank will return the check saying that, sir, there is no funds. What if even if funds there, but they still said there is no funds? Exemplary or vindictive damage. Very good. Now what will holder do? Holder will directly go in auto to the drawer. Ano. Hey, collar idkondo. What did you do? Huh? One payment can't you do? Now you go and threaten him. If at all he is scared of the threatening, he will make the payment. Drawer, payment to be made within 15 days. But no, nothing, no difference. Your threatening did not threaten him. Now what will he do? Holder will directly file a case in the court. Hello. Which court? Not required for us. Don't worry. No, sir, I will go and file a case in the court. The court can order any of this for you. Congratulations. You can go and sit in imprisonment now. You won a jackpot. You have earned a free stay with food. With 100% tight security for 2 years. Is there no life threat at all? No matter what, your life is safe. So with all luxuries and amenities. So people, 2 years you will be imprisoned or up to 2 times of the amount of check. 2 lakh is the check value, 2 times. So 4 lakh rupees can be a fine that can be charged on you. Clear? Huh? This is what this process is called as what? Check bounce. All this is not required for us. Leave it. Clear? Huh? Hello. Hello. என்னடா ப்ராப்ளம் மனசிலாயோ Rules of compensation, huh? What are the rules of compensation? Now see here, machan. Whenever I am getting compensation, that means what? You did not make the payment on time. Then I am getting compensation. Dishonor of bill or note or check or something has happened. So I am getting compensation. For this, there are certain rules, it seems. Now what are the rules? the holder is entitled to the amount due upon the instrument together with the expenses properly incurred in presenting, noting and protesting. What do I mean by that? I will also get the money mentioned on the instrument. How much? 2 lakh. In addition to that, I also will get expenses incurred. Meaning what? Simple lawyer charges I have incurred 1 lakh. I can recover it from you. Hello. Okay, next up. When the person charged resides at a different place from that at which the instrument was payable, the holder is entitled to receive such sum at the current between understood? Sir, now if you look at it, where is the bill payable? Where is it payable? Imperial Bank of Rangoon. Correct? Yes or no? Who should pay it? Somasundaram Jettiar Ano. Correct? Hello. Now Somasundaram Jettiar got a very good package in Google. Now where is he? He is in US. For making your 20,000 payment, he will spend 1 lakh in ticket and come. Then how will he send the money? He will send it through bank. They're telling you how much money is to be sent. You have to calculate in such a way that the day you are sending the money, you take that day's rate of exchange. I need to get 20,000 rupees. Today, $1 is equal to 89 rupees. ಆಯ್ತು ಬಿಡ್ರೋ ಯಾವುದು ಸಾರ್ 87.8 ಸಾರ್ 15 hours questions ಎಲ್ಲ ರಾಂಗ್ ಹೇಳಿ 20,000 now I will divide it by 89 whatever comes what comes maths 100 $1 is equal to 100 rupees see in law we can make anything happen. How much? So people, I need to send $200. Who? Mr. Somasundaram Chettiar. But remember macha, in the transfers there will be commissions involved. All that will be there. So don't be little conjuice. Add another $5. Because who will pay? That should also be paid. Somasundaram Chettiar Anna, you have to pay noda. That's what they're telling you. Understood? Current rate of exchange. That's the meaning of this. Hello?
Yes, sir.
An endorser who, being liable, has paid the amount due on the same is entitled to the amount so paid with interest at the rate of 18% per annum from the date of payment until tender or this understood? No. A, B, C, D. You know this example, huh? You know it, Then okay. Then you guessed it. Who is the next character? See, you know. Hey, you know it. Simply testing. Now you will remember. A has given people promissory note. A has given promissory note to B. Now people, what has B done? B has endorsed it to D. D has endorsed it to C. Now C people has gone asking for payment. A dishonored the bill. Now C went back and took money. C went and of course, whom will C question? Who gave me the bill? D gave me the bill. I went and I questioned D. Yeah, you told me to go and collect the money. That person did not make the payment. Now what do I do? D said, don't worry, I will make the payment. For his self-respect, he paid. Now you tell me, technically, who should make the payment? A dishonored. A did not make the payment. He became insolvent. Now for D, who should make the payment? D also will go and tell the same thing. Hey, you gave the instrument to me. You pay me the money. Now people, B will take some time to pay. It can be immediately. It can be 1 month. It can be 1 year. They are telling you B has to pay whatever is the money you need to pay plus interest at the rate of 18% per annum to the person whoever made the payment. Technically, which is to be paid by you, but for self-respect he paid. You pay him back along with interest of 18% per annum. Understood? Hello. That is what is given here. When the person charged and such endorser reside at different places, the endorser is entitled to receive such sum at the current rate of exchange. Same thing. Now, where is in the same case B and D? Where is B staying? B is staying in US. Where is D staying? D is staying in India. Same continued example. Now, whatever we saw in condition number 2, same thing will apply. Remember, rule 4 is nothing but rule 2 plus rule 3. Hauser, see, rule 3 speaks about endorser. Rule D talks about endorser. Rule 2 talks about current rate of exchange. Rule D talks about current rate of exchange. Understood? Hello? Fifth one, the party entitled to compensation may draw a bill upon the party liable to compensate him payable at sight or on demand for the amount due to him together understood? What is that? Now, sir, D has to get some money. How much he has to get? 20,000 plus 18% interest. Now, what is a guarantee that this B will pay? Now, people, what will D do? Macha, B, do one thing. I don't believe you. You draw me a fresh bill which will include all these expenses put together. We no longer want this bill because on this 100 people are liable. I want you to be liable. Now, B people will draw a fresh bill which will include the original payment plus all the accumulated expenses. Done. Understood? Hello. Nitish Anna. Clear? Pakkana? That is only rules of compensation. Clear? Hello? Done? Okay. So, I think we completed your the business law. So, wish you all the best. Nah? Hey, okay, I'll tell you that. What is that? That 2-3 parts I'll tell you how do we do. So, with regards to exams, as I told you people, business law, try to pay more attention, more focus, write and practice, solve as many questions as possible. That part I will give it to you. And what is that? That tricky questions part I'll give it to you. You can have it, you can study. And to that, if possible, you guys also put more effort from your end. You solve more from your end as well. So make maximum utilization of whatever resources that is already uploaded and available. Yeah. So that is something which I tell you. And yes, all the very best. Do well. May God bless you. Wake up every day, 5 o'clock, whichever God you believe. Spend at least 5 to 6 hours with God. If not, spending on book. I told if you are not spending on book, spend with God. See, something should work. Logic, I am telling you. At least believe in magic. Let something help. What, Pramod? So, chalo people, take it seriously. Do it good. Yes. Thank you so much, people. See you all. Thank you. Same to you. Thank you. Thank you. Oh, congratulations. We did law in 2 days. 3 days, my God. Oh, yes. Thank you. Same here. Miss you too. We'll meet in CA Inter. You'll be there. Hey, I'm healthy, da. Aggressive, da. Of course, I'll be here only. Anything, I'll be roaming around here only. If you come here, if I'm not available, walk to the road end. I'll be drinking tea there. The maximum I'll be here only. So, thank you so much, people. See you all. I hope yesterday you guys have done with your you guys have watched the most important topics, and I hope some topics which you might have left, you have considered it, you have revisited it, you guys have now studied it again, and you are now sitting here. And I know most of you have been waiting for this particular session, that is your detailed case analysis, that is whatever the case laws that is there in our ICAI syllabus I have taken up here. So I will tell you what is the agenda of this. Now in our book, there can be, there are more than, 50, 60 case laws in our book. Some case laws will be very much in detail. For example, if you look at, say, Carlyle versus Carbolic Smoke Bowl Company, the case law is in detail. That is, our syllabus itself, they have given you facts, they would have given you analysis, they would have given you judgment, everything would have been the case in the case of Carlyle versus Carbolic Smoke Bowl Company. But whereas there are some other cases that they would have given one generic line, in the brackets they would have written the name of the case law. Now, the question was, should we consider such cases? Is it important or not? Now, for you, you wouldn't know. They would have given you a line, but they would have just given you that particular case in that particular bracket. Now, we do not know whether that particular thing is important for us or not, and what actually happened in that case law, and when should we quote. So what did I thought is, why don't I make a particular video for all the cases put together, that is everything in your book with background, meaning what happened in short, when this happened, and what was the judgment, and basically what was the rule that was derived out of this case law. So on that thought, this particular case law series came out, and so you can see these are the page numbers that is there in the book, and that is all the cases that is there in our book. So one request for all of you, this is something where I'm trying to work towards on. This particular product is not completely ready. We are trying to do, I'm trying to do something on this particular thing. So meanwhile, please don't ask for this particular thing. So I would be discussing everything, whatever is there. Please watch, the entire thing, but it is not yet ready. If it is there, I would have definitely given it to you. So this is something where I'm not willing to give it in the public domain directly as of now. So please watch, relax, whatever is required from your exam point of view, make best utilization of that part. But yes, please excuse me, wherever it is there, I will only give it to you. Wherever it is not possible, please don't. Please, I hope you guys understand. Yes. So with that, let us start, people. So all the cases have been divided based upon, it has been classified based upon the chapters as well as the units. So yes, let's start with Indian Contract Act. There are some cases where even I am also trying to see what is, because I have to give the complete background and everything. So this is how this particular case law has been done. Okay, yes, people. So let us start. The first one, people, State of Gujarat versus Raman Lal S & Co. You can see here, key principle, meaning what was derived out of this case law. Facts, what happened. Analysis, what the court discussed and that day what happened. Conclusion is, what was the final verdict given by the court. So this is how we are, planning to do. But yes, State of Gujarat versus Raman Lal. In this case, what happened, people? There was ABC partnership. The partnership was getting dissolved. So in the partnership, there will be lot of assets, right? So after the partnership firm gets dissolved, what will happen to the assets? The assets, of course, will be shared amongst all the partners. Don't you think so? So A, B, and C will take those assets. Now what happened? When the assets were getting transferred to the partners, there was an officer, that is a tax officer, IT officer, you can take it as. The income tax officer considered this transfer of assets from the partnership to the partners. He said this will amount to a sale. It's a transfer. and hence as per our tax terminologies, we have to pay tax on it. So Mr. A has to pay tax, B has to pay tax, C has to pay tax on it. Because you are transferring the assets from one person to another. ABC is the person. No, for a partnership firm, you are transferring it to another person. But in this case, it was decided, people, that remember, a partnership firm is never considered as a separate legal person in the eyes of law. From time beginning, from first to second, we will be telling that partners and partnership firm are one and the same. They are not two different individuals. And hence, in this case, a contractor, there has to be two parties. Partnership firm cannot be considered as one party because it is not different from its partners. And based on this grounds, people, this was not considered as a sale. So legal principle, two things you guys can consider here. Separate legal entity. Partnership firm does not have a separate legal entity. Hence, it cannot be considered as a person. And hence, there are no two person in this contract. There is no two person in this transaction. And hence, you cannot have a tax on this. Was what discussed in this particular case law. That is State of Gujarat versus Ramanlal S & Co. Simple. People crazy. Yes. Clear. Okay, that is our first case law. Next one. Balfour versus Balfour. What is a legal principle? The legal principle is, people, legal intention to create or intention to create legal relationship. Husband and wife. Husband had promised to pay some monthly payment like a pension or your allowance every month. The husband had promised wife that I will take care of your monthly allowance by sending you, let us imagine, 5,000 rupees every month. A husband gave a promise to a wife. As promised, husband also gave 5,000 rupees for a period of 3 to 4 months. After that, the husband stopped transferring this money to the wife. Now the question is, people, the wife said, husband had given me a promise that he would transfer 5,000 rupees to me every month, but he stopped transferring. There was a promise that he would transfer 5,000. I gave an acceptance. Now he has stopped transferring and hence he has to transfer it to me. If not, it is a breach of contract. So he stopped. The wife went and filed a case on the husband because he stopped paying the money. Now the question is, people, in front of the court, can I even take up such cases where a husband promises something, a wife promises something? Can I take up such cases in the court? In this case, it was decided that, people, always remember, in case of domestic and social agreements, in between people, they keep exchanging hundreds of promises. Not all the promises they intend to fulfill. Amongst friends, you guys will be promising 100 things. Not everything can be taken up by the court. Now we have to consider these things as domestic or social agreements where you guys do not have an intention to create legal relationship. You never meant to file a case on one another when you guys entered into a contract. And in the court, the case was held in the favor of the husband, saying that, see, not every case the court can take up because these are domestic agreements. Not every promise you were serious. You did not intend to always fulfill all the promises you make. Certain are nonsense, like you guys give it in the class. Sir, this time we are only the toppers, sir. After 10 days, you also won't come. Class only will not come. Forget topper. Now, can I come and file a case on you in that regard? Answer is no. Yeah? So, domestic and social agreements, Balfour versus Balfour. Intention to create legal relationship. The main thing is social arrangements or domestic arrangements. Clear? Done. Lalman Shukla versus Gauri Dutt. What is this? The main thing that happened here is, people, whenever a person asked one person to go and let us imagine this person had a missing dog. I'm just telling you in easy way. I'm not or okay. Again, that also you guys will do on controversy. This person had a missing, let us imagine his son was missing. So what did he say? He went and asked his maid, can you please go and search my missing son? He said, okay sir, anything for you. The maid went and started finding the son. Now, in between this person, the owner was also not sure whether this person will do a good job or not. So, what did he do? He also gave newspaper advertisements. He also printed some flyers saying that anyone who gets my son, I'll give them a reward of 1 lakh rupees. After 2 days, the maid actually found the missing son. So, the maid gave back the son and he went back home. Later in one of the place, he saw an ad that the owner had given an ad. Whoever finds my missing son will be entitled for a reward of 1 lakh. So the maid went for asking for the 1 lakh rupees reward. Now the question is whether the maid will get that 1 lakh rupees reward or not. The answer is yes, the maid will not get the reward. The reason is, remember, yes, you are thinking that, sir, you are cheating. No, people, always read the law as law only. Do not see it with your heart. You have to see it with your brain only. The maid was not aware of the offer at all. Now, in the court, if the maid can prove, I was aware of the offer, yes, the maid will win. But in the court, people, it was proven by the owner that when I told him the condition, the award was not yet decided. So he was not aware of the offer. He agreed to find the missing son even before he was aware of the offer. So he cannot claim the offer. And the legal principle here, people, is always what? It is, remember, the person to claim a contract, to claim an offer has to be communicated. If you are not aware at all, then how can you fight? Yes or no? So, communicated knowledge of the offer is important. If that is only not known, you cannot fight. That is a case law done. Harvey versus Facey. What is Harvey versus Facey? Also called as bumper hall pen case. Simple. One person liked another person's land. The land is called as people bumper hall pen. In various places they would have sent pen means pen. It's not pen, people. Bumper hall pen is a name given to a house. So one person wrote a letter to another person. Would you be interested to sell your building to me? So this person replied, people, he said, would you sell your land to me, meaning building to me, and what will be the best possible price that you would be selling your land for? This person, so there were two questions. Will you sell your land? Next one, people, what will be the best possible price? He just replied for the second question, the best possible price is 900 pounds. I replied 900 pounds. That's the best possible price. Now, A replied, I'm okay with the price. Thank you so much. When can I come and collect the keys? This person replied, I never wanted to sell you. You asked me what is the price. I said 900 is the best possible price. He said, no. I clearly said if you are interested, you have to say what is the price. When you said price, that means you are giving your acceptance. So he started fighting for it. In this case, it was decided, people. Remember, when there are clearly two questions asked, just giving a price does not amount to an acceptance. So mere quotation of a price is not a contract. It does not amount to an offer. It does not amount to an acceptance. A clear yes or a no should be there. Just me telling a price cannot be considered as acceptance. Harvey versus Facey. Yes. So no contract arises unless a clear offer is made and accepted. Mere quotation of a price is not an acceptance. That is the main principle you need to write. Is this clear? Cut, copy, paste cases. Macpherson versus Appenda. Cut, copy, paste. See, as in Harvey versus Facey, same thing happened here. The owner of a house stated that he would not accept less than 6,000 euros. So same thing, I wanted to sell my land. The other person said, what is the best possible price? This person said that I will not accept anything less than 6,000. So the other person said, then okay, I'm okay with 6,000. I said I will not accept anything less than 6,000 doesn't mean that I'm okay to sell at 6,000. I said if someday something comes, I will not go for less than 6,000. So these things cannot be considered as an offer. It has to be clearly communicated. No contract arises until offer is made and accepted. Same, cut, copy, paste. Now sir, people, you guys would be having a confusion. Should we follow Harvey versus Facey or Macpherson versus Appanna? Which one should we follow? Facts are same, scenarios are same, conclusion is same. You can ignore this. That's why in our books we would have popularly followed Harvey versus Facey. That's the logic. Understood? Okay, done. What is this? Harris versus Nickerson. An auctioneer advertised that certain goods would be sold at an auction. The plaintiff traveled to attend the sale, but the goods were withdrawn. See what happened? I've given an advertisement in a newspaper that the auction will take place from 10th of September to imagine 13th of September. There is an auction. So one person came all the way from Delhi to participate in this auction. But people, the auction was finally withdrawn. On 10th people, there was no auction held. So the person filed a case on the person that there was an offer and this person did not, what does that say? But the goods were withdrawn. Or you can take it like this. Imagine on 10th of September, I wanted to sell 10 items. In that I sold only 8 items. 2 items I did not sell. So a person who came to participate in this auction, he came for those 2 items only by looking at an advertisement. But the question was people whether is this person liable for that person. First of all, people always remember, I hope now your mind is running, how to write the case laws. Yes, people, as you guys rightly said, the case law will come. What? It is just an invitation to an offer. We are calling you to participate in the auction. I am nowhere liable to the articles now. I have told I will be selling it. Can I recall it? Yes, revocation of an offer can be done before acceptance. It is my choice. Are you getting the point? See, I gave an invitation to an offer. Just by coming here, is it an acceptance? No. In the invitation, in the bidding, if at all you want the highest bid, then the acceptance will come into picture. I hope this is clear, all of you. Understood? That is what was held in Harris versus Nickerson. So withdrawal does not amount to any breach of contract because a contract has not yet come. A tender, advertisement to a tender is just an invitation to an offer. Simple. Boulton versus Jones. What is the principle? Specific offer, specific acceptance. A specific offer can be accepted by a person to whom it is made. A gave an offer to B. So B owns a shop. A said I wanted certain items and he wrote a letter to B. Can you please sell these items to me? B sold his shop to C. So next day morning C opened the shop. So C saw the letter written by A to B. So it is his shop now. So C sent the goods to A. Now C after 2 days asked for money with A. A said I will not be liable to pay because there was certain dealings between A and B. There was certain dealings with us. Why did you come in between? Now the question is people, can C recover money from A? Answer is no. Because this is considered as specific offer. When A has clearly written an offer to B, it is B's responsibility and not C's responsibility. Specific offer can be accepted only by a person to whom it is made. Boulton versus Jones. But remember, C has a right to recover the money from B. Always in your classes, when you guys are reading, you always will have this confusion. Sir, then Papa knows Sir C. People, I'm not saying that this person will not get money at all. He will of course file a case on B. He will recover the money. But not from A. A is nowhere relevant. Because with them they had some other private dealing. Are you getting the point? All of you? 100%? Case law Boulton versus Jones. Specific person cannot be accepted by someone else. An offer made to a specific person cannot be accepted by someone else. Done up. Next one, Carlyle versus Carbolic Smoke Ball Company. A general offer, open offer can be accepted by any person, public at large. Anyone can accept it. And remember, acceptance need not be communicated. Following the instructions given in the advertisement itself will be considered as an acceptance. In this case, what happened? There was a company who gave an advertisement in a newspaper that if at all anyone who uses our medicine and if you still end up getting up that time, there was something called as influenza like COVID. Imagine, I will tell you like today's scenario. If a company comes and says you take our tablets like a immunity tablet, even after taking, if you get COVID, then they are telling you that we will be responsible. You will be eligible for a reward of 1 lakh rupees. So there is an innocent buyer who goes and purchases those medicine, who takes the tablets as per the instructions given. One in the morning, one in the night. He took it for 20 days. After taking also people, this person ended up getting COVID. Will he have any right? Answer is yes. This is called as what people general offer. General offer means when you give a newspaper advertisement, whoever reads it and who acts upon it will be eligible to get that particular benefit. Remember the difference between this and Lalman Shukla versus Gauri Dutt. In this person was aware of the offer. In that he was not aware. And you acting as per the instruction. What is the instruction here? Take 2 tablets, one in the morning, one in the night. That itself is an acceptance. It need not be communicated. That is Carlyle versus Carbolic Smoke Ball Company. Is this clear? Done. General offer. Next one, people, Neil versus Merit. What does that, people? Always remember, rules of acceptance says that the acceptance has to be unqualified. Meaning what, people? The acceptance should not have any conditions attached. Meaning what, sir? If at all I am saying, I want to sell, A wants to sell his car. In this case only I will tell you, A wants to sell his car to B. At what price? A wanted to sell it for rupees 5 lakh. Now what did B say? B said, yes, I am okay with it. He also gave 1 lakh rupees as an advance check. And he wrote a letter saying that the rest of the 4 lakhs I will give you in 2 installments of 2 lakh each. I will repay it within next 2 months. Is it okay? So 5 lakh I have agreed. But I am telling 1 lakh I will give you now, 2 lakh I will give you next 2 months. Now is this a valid acceptance? Yes, you guys rightly said it is not a valid acceptance. Why? Why na? Because think. Because I just said I want 5 lakh. Did I ever mention you that you can give me 1 lakh now, another 2 lakhs next month? Did I ever tell that? No. So this is what is called what? Conditional. This becomes what? Counter offer. Qualified acceptance is always counter offer. Now you are saying I will buy your car provided if it is sold in EMI. I should be okay with it. Now yours become offer. I should give an acceptance. That is this case law. Qualified acceptance is never a valid acceptance. Acceptance should always be unqualified, unconditional. That is the word. So these are the provisions. If you find such things in your book, in the question if these stories are coming, then you have to quote these things as valid case laws. So when we are writing our exam, I told you last day in our Mission 80, I told you that I will tell you how to present your answers. In that I will show you how to present when we have similar case laws. Clear? Okay, done. Now, what is this? Counter offer. Union of India versus Bahula. In this case, what happened, people? A wrote a letter to B. A wanted to sell the land. I asked, let us imagine. A wrote a letter to B saying that I want to sell my land for 30 lakh. Are you interested to buy? B replied, people, yes, I am interested to buy, provided if you sell it to me for 24 lakhs, I will buy. Now, of course, this is called as counter offer, conditional acceptance, negotiation. So the first offer came to an end. So always first offer comes to an end. Now it is A who has to give an acceptance, whether I am okay with 24 lakh or not. Now in this case, what happened, people? A was not okay with 24 lakh. Now B later on, after 2 days, said, okay, I'm okay with your initial offer that I will buy it for 30 lakh only. Now the question is, people, is this a valid acceptance? Now is this a valid contract? That was the question. Yes, people, this is a little tricky. The answer is it is not a valid acceptance because when a counter offer was made, the first offer came to an end. The first offer is done. There is no longer that is existing. Because of your counter offer, that offer came to an end. Now your 30 lakh itself will become a new offer. Now A will have to say yes to it. That is this case law, Union of India versus Bahulal. What does it say here? Once an offer is rejected or a counter offer is made, the original offer cannot be revived. The same thing cannot come back except by the offerer. No contract exists until the offerer accepts the counter offer. Now A has to accept that. Here all of you. Yes, nice one. Next one, Brompton versus Metropolitan Railway Company. Same thing, people. This is opposite to Lalman Shukla case. What is that? In Lalman Shukla, offer has to be communicated. In this, people, acceptance has to be communicated. A simple thing, a company wanted to approve a certain company as their raw material vendor. Let us imagine there is a company A. We wanted to give a contract to a person, that is B, to supply raw materials to us. So company B gave us a quotation that this is what will be the price. So in company A, there was a manager. The manager saw the quotation and he wrote approved and he kept it in his drawer. Now the question was, offer was made that raw material 1 kg will cost me 1000 rupees. I said I'm okay with it. I approved it. But where did I keep it? I kept it in my drawer. I never gave it back to Mr. B. Now the question is the contract coming into picture? Is the contract existing between A and B? Yes, as you guys rightly said, there is no contract between them. Why? Logically think. B does not know what you did with that paper. Allah, you wrote approved, you went and took Bel Puri, Anna, you ate something. How do I know what you did with that paper? Understood? Acceptance must be communicated. Brompton versus Metropolitan Railway Company. Done. What all names are coming? Okay. Sir, Bhagwan Das, Govardhan Das, Kedia versus Girdarilal, Parshottam Das and Co. My God. 1966. In this case, what happened, people? The appellant, now see, it's a nice, different one. People, now see, if you see all these cases now in our book, we will not have complete facts. But because the case is there, a scenario may come. So that's why I thought, okay, because the words are there, let us look into the case and let me explain you at least in short. Now when they are asking you, remember this, okay, it is something there. And from your end, at least put little effort. See, I have paused it for a while. You can take a picture, you can take anything that. Take a minute to write a note, please. Yes, can you guys do it? Please, show me your cooperation. Say cheese. Very good. Achhe pyare bache. People, okay, in this case, what happened, people? See here. Whenever, see, the contracts can happen in 3 ways. One is when people are standing right next to each other, easiest way of contract. Next one is by posts. Third one is by telephone. So in a telephone contract, what will be considered as place of contract? Like, let us imagine a person from, if you guys remember in most important topics, I have given this also. A is in Bangalore. I'll take the same example I was given in most important topics. A is in Bangalore. B is in, I think I have taken Hyderabad. B is in Hyderabad. A gave a call to B, I want to sell my car for 5 lakh, are you interested? B said, yes, I am interested, I will buy your car for 5 lakh rupees. Now this, the question is, what is considered as the place of contract? Is it Bangalore or Hyderabad? Why is it important? Tomorrow, imagine if there is any dispute between you guys. Where will you guys go and fight? Is it in Bangalore's courts or will you guys go and fight it in Hyderabad's court? Where will you go and fight? In this case, it was decided wherever acceptance is received will be considered as the place or the jurisdiction of that particular contract. Now, where is acceptance received? Acceptance is received wherever A hears yes, I am interested. So, in Bangalore, I am hearing correct? That is what they are telling you. The respondent accepted. When the appellant failed to take delivery, the respondent should. The telephone conversation is instantaneous form of communication. Unlike postal communication, acceptance is effective when and where it is heard by the offerer. Therefore, the contract was concluded in Ahmedabad and the courts there had jurisdiction. So, Ahmedabad here is in our case is Bangalore. See, complete when the acceptance is heard. Clear, all of you? Pakka. So, wherever I hear the acceptance will be considered as a jurisdiction of that particular contract. Done. Simple case law. Done. Next one. What is it? Hayworth versus Knight. This is not a very good one. We do not have much in detail. This is nothing but people, minor variations in the wording of an acceptance that do not change the substance of the offer, do not invalidate the acceptance. What do you mean by that, people? Now imagine, people, I am selling you my car for 5 lakh rupees. I am telling you, I want to sell my car to you for 5 lakh rupees. Now you reply to me saying that, people, I want to buy your car for 5 lakh rupees as told by you. Now what is that? I am not actually accepting in the same words as you said. I might be adding 1 or 2 words here and there, but the meaning is not changing. Meaning I am not adding any conditions to it. Sir, did not understand. Meaning, your exams are, they are expecting you to write what is voidable contract. What will you write? Voidable contract means a contract which is valid or invalid. Correct? Meaning is same. But what are you expected to write? A contract which is voidable at the option of one party but not at the option of other. Meaning is same. Intention is same. But the way you are communicating is different. They are telling you in this case, as long as the intention is same, the words, if at all here and there 1 or 2 words are getting added, that will not amount to cancellation of a contract. It will still be a valid offer. It will still be a valid acceptance. But I am not telling you it should be variation. Variation means it will become qualified acceptance. Wordings can be different. It is okay is what was discussed in this particular case law. Not so important. Okay. If you are planning to remember so many cases what to do, this is okay. You can leave it. Next one, Feldhaus versus Bindley. What is Feldhaus versus Bindley? Silence cannot be considered as acceptance. A told B that I want to buy your car. If I do not listen anything back from you, I will consider it as an acceptance. So such things cannot be valid acceptance. Acceptance has to be either orally, written or by conduct. You should say something. Sir, the offer cannot have a term that if you do not accept, I will assume that you are accepting it. So that is what was discussed in this Feldhaus versus Bindley. Same thing in the case car put horse. So one person said, if you do not say anything, then I am assuming that you are interested to sell your horse to me. It cannot be considered as valid acceptance. Next one. I hope you guys are understanding that. Hey, let me know. Central Bank of India, Yacht Mall versus Venkatesh. Mental assent or uncommunicated resolution does not amount to acceptance. Acceptance must be communicated to the offeree. Same thing. A bank resolved to sell land to A but failed to communicate its decision. The court held that merely passing a resolution did not create any contractual obligation since the resolution was never communicated. Meaning what? Imagine in a bank auction, one person had taken a loan and he had taken a loan on a property, and this person does not repay the loan. Now what does the bank decide to do? The bank decided to sell that property in an auction, and they decided also in the bank, they passed the resolution. Let us sell off this particular product. Let us sell off this particular product. This is more clear. This is more clear. Hello. This is clear? Yes. So the bank passed the resolution also that let us sell off this property, but it was never communicated to the other party. So same thing was discussed and decided in this case law also. As long as it is not communicated, you cannot assume that there is a contract. Always it has to be communicated. Acceptance should always be communicated. Here. Okay. Planning to remember, you can leave it. Enters Limited versus Miles Far East Corporation. Cut, copy, paste whatever was discussed in the case law of Bhagwan Das Govardhan Das Kedia. In this case, what was decided? Whenever instantaneous contracts, meaning what people, whenever it is over telephone, wherever you receive will be the place of contract. Cut, copy, paste is this. Nothing will change. Can you see this? Clear? Same? Done. Mukul Datta versus Indian Airlines. What is this, people? Nothing but special conditions. People, for this we would have seen this case law in our class. Lily White versus Manuswamy. What is this case? Remember, people, whenever in a contract, you'd be entering so many contracts, right? Like for example, I want to travel in a flight. Now, behind the flight ticket, of course, now everything is electronic, things are changing. But at least if I go back 5 years, I used to get electronic tickets. I used to get physical tickets. Now the question is, whatever is given in the tickets, you guys would have never read it. Are those conditions binding upon me? Does it bind me? I have not read it. Will it bind me? The answer is so will it bind me? That was a question, right? Will it bind me? The answer is, people, always remember, if the conditions printed on the tickets or any place, you go to a movie, you go to a shop, you're getting an invoice. If the conditions are reasonable, then it is binding you whether you have read it or not. And that is what is considered as special conditions. So if I have to combine Mukul Datta versus Indian Airlines and Lily White versus Manuswamy, the verdict, conclusion is same. If there are any special conditions printed on a ticket and if they are reasonable, then it will bind the parties. Exactly that was discussed in Mukul Datta versus Indian Airlines. So a person was traveling in a the aeroplane. So in that, whatever tickets, he said there are some conditions. After everything happened, that this person said, I did not know. The aeroplane said, of course, you guys, it is printed on the ticket, you are liable. It was discussed finally in the court. It was decided that if it is printed on a ticket, you are liable. There is no going back. In Lily White versus Manuswamy, other way around. It was printed. One lady gave her sari for a laundry. The laundry people ended up missing that sari, but on the ticket it is written, if at all we miss your sari, if we make your product unfit, or if we make your product unusable, in such cases you will be entitled for a compensation at the rate of 15% of today's market price. Whatever is the value of that product today, in that 15% will give it to you as compensation. In this case, court decided and said, special conditions people, if at all it is unreasonable, then it will not bind you guys. Then you need to claim something more as compensation. So special conditions, but if it is not, valid, if it is not reasonable, then it will not bind the parties, was what discussed and decided in Lily White versus Anuswamy. Okay, what is this? What is this? Raipur Transport Company versus Ganesha. What is that, people? Okay, imagine like this, people. ArivuPro sells our classes to the students. I don't know if I can give this example or not, but we shouldn't actually. But yes, for you to understand better, I'm telling you. ArivuPro, we sell our class to the students. Meaning what? Let us imagine I take admissions for CA Foundation and CA Inter. Now we have clearly told people while we are giving you an admission, people, if you miss classes, if you miss attending the classes, you guys will get the access for recorded videos. If you miss also, you need not worry. You can still watch it on a recorded content. Now, what will students start doing? Here and there, they will start missing the classes wantedly without reason. They will end up piling the syllabus so much that they can't watch recorded videos also. Now, what will ArivuPro do? After you guys join, now sale has happened. We said if you miss, you can watch recorded videos. After you guys have purchased, you have come to the classes, you have sat, on day first, on orientation, we will tell you. So now what I'll do, once again, some problem. So now what we will do on day one, orientation, what we will do, I'll only tell, if you guys miss classes without proper reason, we will say, if 60% minimum attendance is not maintained, we will not give you recorded access at all. Now the question is, people, is this condition binding on you guys, on students? Can they say that no, it is not binding, or can we say, hey, it is our discretion, we can impose any condition? The answer is, people, technically, don't tell to anyone. Yeah. People, and don't tell management I told this, example purpose I'm telling you. People, this will come under conditions imposed after contract will not bind the parties. After the contract is made, if at all you want to enter into any new terms and conditions, it has to be always with mutual agreement. So this can we do? Answer is no, is what was decided in this case law. Special conditions inserted after a contract is formed are not binding. Pakka, what this case law is. Done. Okay. Next one, sir. Ramsgate Victoria Hotel Company versus Montefiore. What is this case law, sir? Okay, in short, I'll tell you. There is a person called Mr. A and there's a company called Ramsgate Victoria Hotel. Victoria Hotel people, they came up with, let us imagine, something called as IPO. They wanted to sell their shares to the public. One of the person, yes, people. So, now in this case, what happened? There is a person who applied for IPO. Say, for example, on 1st Jan 2026, he applied. The company never allotted the share to this person. Allotment meaning the acceptance was not given. So, now in this case, the question is, people, on 1st Jan he applied. Even by end of Jan, they did not give allotment. End of Feb, they did not give allotment. End of March, they did not give allotment. So, this person thought, people, it is done. But somewhere in the month of June, yes, people, we were doing this case law of Ramsgate Victoria Hotel Company versus Montefiore. In this case, what happened, as I told you, a person applied for an IPO on 1st Jan 2026. The company did not give an allotment even on 1st of Feb, 1st of March, the allotment was not given.
Now the question is, people, whether okay, in until 1st of March also it was not given. Now what did the company do in the month of June when the market price is down? So imagine if the face value is 10 rupees, the market price that time has become 5 rupees. That time, people, they gave allotment to this person. Now this person is rejecting the offer, saying that you cannot give an allotment after 6 months after IPO has come into picture. Now the question is this valid acceptance by the company or not? They gave an acceptance in the month of June. So in this case, it was decided, people, acceptance must be communicated within reasonable time. So whatever the IPO allotment the company gave in the month of June is not considered as reasonable time. A month or 2 maximum can be considered as reasonable time, but not 6 months or 1 year cannot be considered as reasonable time. Cut, copy, paste, Ramsgate Victoria as well as Indian Cooperative Navigation and Trading Company Limited versus Padam Se Premji. Cut, copy, paste. Yes, allotment was invalid because it was made after unreasonable delay. Simple, done. Next one, sir, unit 2. What is this? Unit 2. This is nothing but, people, Misa versus Curie. In this case, it was held, people, consideration can be a positive act as well as a negative act. That is, it can be to do something or abstain to do something. That is what was this case law. So, someone said, I will give you money to discharge the debt of a person, was also considered as valid consideration only. Exam point of view, I would say still okay, but what is the main point here? Abstain. That is, it can be positive as well as negative. That was the main verdict of this particular case law. Till now, people, I was sitting up, we were doing no, this is proper Ganesha mantra. We speak, 100 speakers will come and say Tamte Dankanaka. So, that is only going on, but yes. Yes. So, after that only we started, but yes. Okay. How much of inconvenience, no? It is good as well as bad. Now right in front of our academy, one road is there. Complete road is blocked. So, in my childhood also, we also used to do, I'm not saying no. But the population then was different. Today's population is different. So much of inconvenience will be caused. But yes. Next one, people. Durga Prasad versus Baldio. What is that, people? Consideration must move always at the desire of the promisor. A told B to construct certain shops. A told B to construct certain shops in a particular city. B constructed those shops as well. Now, A told B, you construct shops in the city and you charge rent for it. Now, B started charging 2 rents. One is to use the place, 1 rent. Next one, he constructed the shop for them. No, he started selling another, a percentage as commission. Because I've spent so much of money, no. For you guys, I've done it, no. So for that, you pay me an extra on your sales. You pay a particular percentage as commission to me. So one is rent and one is commission. Until one day, people, where one person came and said, why should we pay you commission? Did we ask you to build? So a person, C, who is taking the shop on rent is coming and saying, did we ask you to build? Rent we will pay because we are using it. Why should we pay this? In the code, it was decided, people, consideration should always move at the desire of the promisor. C never asked you to build the shop. So you cannot claim for construction also you have to pay a particular rent. That is not allowed. That is not binding on the other parties because they never asked for it. Durga Prasad versus Baldio. The key principle is, people, what? The consideration must move at the desire of the promisor. Done. Chinnaya versus Ramaya. Consideration may move from the promisee or any other person. A old lady said, I will give you my properties. All my properties, I'll give it to you. Chinnaya said to Ramaya that I'll give you all my properties. I have only one condition, that I have one brother. You have to give him every month some pension for his monthly living. She said, okay, I will give. After promising, people, she said, this old lady passed away. They gave the property and passed away. But Ramaya said, going forward, I will not give you even 1 rupee because I am giving you pension. What are you giving me? There is no quid pro quo. But in this case, Chennai said, whatever my sister gave, that will be a consideration on behalf of me. So consideration may move from promisee only or any other person. It will be a valid consideration. This is clear. That is what was decided in this particular case law. Next one, Kedarnath versus Gori Mohammed. So in this case, what happened, people? I think I told you in the most important topics also. What is charity? You agreeing to give. Imagine Mr. A saw one advertisement on Instagram that one particular child is suffering from cancer. So A said, I will give, he messaged, I will agree to donate 10,000 rupees towards this particular patient. So like that, lot of people started doing it. So the people who were collecting the donation, they decided to go and admit that child to a hospital and they wanted to get the treatment done. Now this person saw the treatment. He saw that, okay, everyone have already given money. Lot of people have agreed to give money. Now why should I give 10,000 rupees? He wants to back out. Now the question is, in a charity, will it bind you or will it be considered as a valid contract? Remember people, in a charity, depending upon your word, if someone has undertaken the liability, meaning they started the operation, they started the surgery, now people, you will be bound by it. You will have to pay whatever you have agreed to pay. So a charity, upon a liability being undertaken, will become a valid contract. You are bound by it. Kedarnath versus Gori Mohammed. Charity is the main principle. Okay, done. Unit 3, Mohari Bibi versus Dharmodas Ghosh. Most popular case law. A child went and borrowed a loan from a major. He was a minor and the contract was considered as void agreement. And what was the verdict? A minor agreement will never be a valid contract. The courts will never help you at all. So the minor will be free from all the debts. But remember, there is also called as something doctrine of equity. Under this, yes, we will not protect. But if the minor has taken 20,000, if the money is there in the bank account, people, under the doctrine of equity, the courts will always tell the minor to return that money. But what if he has spent? If he has spent means people, then karma. We can't do anything. But if the money is available, the court will always recover it for the person. Because we cannot make a misuse out of the law. Clear? Mohari Bibi versus Dharmodas Ghosh. Sain Das versus Ramchand. What is that, sir? In this case, there was one major and there was one minor. Together, they borrowed one loan. Whenever there is a joint agreement in which there is one major, one minor, minor will not be liable, but major will be liable. Joint promisors where minor and major both are involved. Minor will be free from liability. Major will be liable for the entire liability. Sain Das versus Ramchand. Key principle, minor agreements. Major will be liable in a joint contract. Clear, Ada? Okay. Next one. State of Bombay versus RMD. Chamar Baugwala. Now in this case, what happens, sir? Simple people, nothing but wager. Crossword puzzle. Is it considered as wager or not? Simple people, if a winner is decided based upon luck, then people, it's a wager. If a winner is decided based upon skill, then people, it is considered as valid agreement. Provided, yes, the prize money does not exceed that 1,000 rupees thing and all will come. But yes, remember that. That is the solution which was decided. It was decided in State of Bombay versus RMD Chamar Baugwala. Simple crossword puzzle. Wagering is the key principle. Are you understanding, Ada? Hello. Done. Next one, Gibbons versus Westminster Bank Limited. In this case, what happened, people? I have told this even in your most important topic also. Remember, people, there is something called as vindictive damage or exemplary damage. It is always awarded whenever you fail to marry a person or whenever there is a wrongful dishonor of a check. Meaning, my account has balance, but the bank wrongfully said there is no money in my account. Now, whose account is this? Is this a businessman or this person is a non-businessman? If you are a businessman, people, by default, you will be entitled for exemplary damage. Revenge you will by default get. But if you are a non-businessman, people, you need to prove what did it affect and how did this wrongful dishonor affect your status. If you cannot prove, then by default, people, we will not be entitled for exemplary damage. By default, we will be entitled for nominal damage. Because there is no effect because of whatever dishonor it happened. We did not suffer any loss. So that's the judgment we take from this. This is clear. Gibbons versus Westminster Bank. Rochester versus De La Torre. What happened in this case law? There is a person called as A. He called B and he said, imagine this person is coming from France and this person is in India. He said, I'll be visiting India in the month of 1st June 2026. Can you be my tour guide from 1st June 26 to 1st September 2026? This person said, okay, I'll be, and they entered into a contract. This person called him on 25th May 2026 and said, I would want to cancel my contract. Meaning I don't want to go ahead. I would want to go back. Now the question is this considered as breach of contract? Because now this person is telling the contract has not started at all. The contract will start on 1st June 2026. It has not started at all. So people, remember, this is called as executory contract. You guys have agreed. Contract is made. Whether it has started or not, it is irrelevant. But you guys have agreed. So it is a breach of contract. So this tour guide will be entitled for compensation. This is an anticipatory breach of contract. Whether will I be entitled for compensation? Answer is yes, I'll be entitled for compensation. Anticipatory breach of contract. I will be entitled for compensation. Done. Next one, Frost versus Knight. Same thing. A promised B that after this person's father dies, I will marry you. He promised. But what did this person do? As long as his father was alive, he ended up marrying another lady. He married another lady. So it is so evident that people, I cannot marry her immediately now. So the law considered this as, again people, a breach of contract by conduct. You entered into a scenario in such a way that now you cannot marry her. You need not have to tell it. We know it by conduct. So now what she can do? If she wants, she can wait. It is left to her. Or can she file a case? Yes. What will she get? She will get exemplary damage. Frost versus Knight. A person promised to marry, she will get a compensation because of a breach of contract by conduct. Here, damages, exemplary damage. That's the case law. Shamlal versus State of UP. We have seen this also. What happened in this case law, people? The case is for a quasi-contract. Basically, what happened in this case law? Okay, so this person was working for one of the government. The government removed him from the job. He went to the court and got a stay order, interim order, that I should not be removed because there should be a hearing. The court also passed an order in the favor of this person. Yes, without hearing, you cannot remove that person. So the government took this person back into the job. So because he was taken back into the job, the government had to pay him salary every month. So they paid him salary for 6 months. Of course, simultaneously, the court case was still happening. The government was sure that it is going to win. The government did not allot even one single work to him in the 6 months. Now after 6 months happened, people, government won the case. The case went in the favor of the government and it was decided that yes, you can remove that employee because of these grounds. The government removed him and the government filed a case to recover this money. under quasi contract, and no one can take a benefit of something which he is not entitled to. 6 months you did not work and you were also aware of it. So because of this, it was decided that this person, Shamlal, has to return the money whatever he has taken as remuneration for which he has not worked at all. That is his case law. Done. Holland versus Howler. What is this, sir? Nothing but people, finder of lost goods. A person went to a hotel. This person saw a diamond ring. He searched for a owner he could not find. So he went and he gave the ring to a cashier. He said someone has lost it. So if someone comes asking for the ring, please give this ring back to them. So after 1 week, people, this person again came. A came and asked B, did you find the owner? Were you able to return the ring to them? The cashier said, no, we were not able to return because no one came in search of it. Now the question is, whom will this diamond ring belong to? A or B? Because the owner is not there. Remember, people, in this case it was decided whoever finds the product will be considered as the next owner. So A found the product. So whatever, let us imagine if this cashier has, spent some money to find the owner, like giving an advertisement or whatever. If he has spent some money, A will have to return that money to B and A can keep the product with him. Whoever found the product will be the next owner. But yes, you need to make sure when the owner comes, you need to return the product. Here are Holland versus Howler. All easy case laws, Noda. Hello. Shri Shiba Prasad Singh versus Maharaja Shrish Chandra Nandi. In this case, what happened, people? In this case, it was decided nothing but people. The case is again revolving around something called as mistake. The royalties were paid under a lease after a lease. In short, people, nothing but remember, if at all any money is paid by mistake, you will see this under quasi contract only. If there is any money paid by mistake, whether it is mistake of law or if it is mistake of fact, any money paid by mistake, whether mistake of law or mistake of fact, that money is still recoverable under quasi contract is what was decided in this case law. Exam point of view, okay, not that important, you can ignore. Sales tax officer versus Banaras versus Kanhaiya Lal Mukund Lal Saraf. In this case, what happened, sir? Same thing again. See, taxes collected under an invalid statute paid by mistake of law must be refunded. Meaning, in short, I'll tell you, people, A did a transaction. Let us imagine he entered into one contract. He did a transaction. There was a sales tax officer who said, this particular transaction will be levied a tax. There is a tax you need to pay. This person paid the tax also. But he said, how am I responsible to pay this tax? This does not come under that scenario at all. But the sales tax officer did not live, so the tax was collected. Later on, it was proved that people, for this transaction, the tax is not attracted at all. I need not pay. But the sales tax officer is telling, no, it was paid by mistake. And hence, next time you need not pay, but for this time it is valid, we will not refund you the money. The law was decided in the favor of this person. Of course, today, what is this exploitation? The law decided that no, whether paid under mistake of fact or mistake of law, money is refundable. Quasi contract, yes, done. Next one, Seth Kanjelek versus National Bank of India. Again, people, what is this? Someone forced a person to pay money. So can I return it? Yes, people, under the words coercion. In this case, what was discussed was coercion includes a lot of things like extortion. What is extortion? Someone blackmailing you to pay the money. Even that is also considered as not valid. If at all someone has taken money from you like that, that can be returned, refunded, quasi contract only. Exam point of view, okay. Trikamdars versus Bombay Municipal Corporation, a person who pays penalty under duress or threat of prosecution. Again, in this case, what was decided is, people, let us imagine I'm going in a bus. I did not buy a ticket. Now a TC comes, the ticket collector comes and he says that where is your ticket? I said I did not buy. And the person says you need to pay a penalty. Penalty of how much, people? I need to pay a penalty of, let us imagine, 10,000 rupees. Yeah. I said I don't have money now. He said if you don't pay money now, I'm going to put you in jail for 2-3 years. He said, sir, I understand I did not pay ticket. I did not buy the ticket. But I need some time to pay this. You can't say that if I don't pay now, I'll be put in jail and all. He said, no, nothing doing. If you do not pay the money now, then I am going to arrest you. Now people, this person called so many people, he took so much of help and he tried to clear that 10,000. And after paying that 10,000, he filed a case against this collector, that is ticket collector, saying that the money was taken by him by force. He was not given a fair chance to pay the money. The money was taken by him by force. They did not give him a fair opportunity to pay. So this money, whatever was taken, was it valid or invalid? People, you will not believe, in this case it was decided that whatever the ticket collector did was invalid. Because you have to say that yes, you need to pay penalty. But remember people, penalties, whichever law, it will always come with a time period. And no one will be moving with 10,000 rupees in pocket. Of course. Now why is this coming under coercion? This was also considered as coercion, you know. And the money was returned. The TC was suggested to return the money collected as penalty because it was not conducted fairly. Yeah, because even that is the duress, the pressure that you put is still considered as coercion. And it was decided in this case that you have to return the money. Logic understood, no, penalty is valid. I'm not saying penalty is invalid. But you need to give certain time period to collect the money. You cannot say that pay tomorrow, is what was decided in this case law. So with the fear of getting imprisoned, he paid immediately, can be returned back. Next one. Gajan Moreshwar versus Moreshwar Madan. Indemnity holder can sue the indemnifier. Meaning what, people? In this case, again, not so important. Meaning, imagine I've taken some insurance. I can ask money from my insurance company as and when I meet with an accident. As and when my bike meets with an accident. So whenever the liability arises, I need not have paid the money. I need not have got it repaired yet. But as and when the liability arises, I can go and I can ask my insurance company to pay me the money. So the indemnifier will be liable to pay the money to indemnity holder as and when the liability arises. Yes, sir. Not when the loss actually occurs, meaning I need not have paid. Liability happens, you will be liable. Done. State Bank of Saurashtra versus Chitranjan Ranganathan Raja. What happened in this case law, people? A principal debtor borrowed money from a bank. He took loan. And of course, bank also took something as collateral, that is security, pledge. Let us imagine gold. And there was also a there was also a surety. The bank, due to its negligence, people, they lost this security. So in this case, it was decided that the surety's liability will reduce by the extent the bank has collected that particular collateral. So imagine if the loan was 1 lakh. The bank lost a gold worth 50,000. The surety's liability will also be reduced by 50,000. Always remember, the surety's liability is coextensive with the principal debtor. And surety has a right over the security interest created by the principal debtor. So surety's responsibility will be to pay 50,000 only. Is this clear? Done. Hyman and wife versus Nee and Sons. In this case, what happened, people? Whenever the case is on bailment, and what type of bailment? Bailment is non-gratuitous bailment, also called as bailment for hire. In this case, what happened? A particular person took, let us imagine in today's scenario, a person took a Zoom car on rent. The Zoom car brakes were not working properly. So the question is, people, a person went and hit someone, so there is a liability. Is Zoom car liable? The Zoom car was not aware that the brakes were not working. So remember, in a non-gratuitous bailment, meaning whenever the money is involved, you have taken it for rent, the person will be liable for all the defects, whether known to him or not known to him. So Zoom car, whether they are aware of that there are defects in the car or not, Zoom car will be liable. Principal non-gratuitous bailment, that is bailment for hire. You will be liable for all the defects, whether known to you or not known to you. That's the conclusion. I hope you're able to understand. Great Northern Railway Company versus LEP Transport and Depository Limited. In this case, what happens, sir? Now imagine people, there is a person, he sent certain goods via ship. So there was a certain goods sent by this person via ship. So like a consignment, you send, no, imagine some export is happening. Now people, this is a bailment, of course. Now, whenever you are bailing people, whenever you are giving certain goods on bailment, it is your duty to disclose if it is any dangerous or hazardous. This person did not disclose the nature of the goods. So the goods were kept in a normal way, that will be kept in a ship. But after it is being kept, people, it was known to the captain after everything was done that there were certain dangerous goods that were kept, because of which the goods around it has been spoiled, destroyed. It was held that the bailer will be responsible because it is your duty to disclose the dangerous nature of the goods. So whatever is the nature of the goods, you need to disclose as a bailer, is the case law. Done. Shantilal versus Tara Chand Madanna Gopalji. What happened in this case? In this case, people, simple. A person gave, imagine this person had some 50 bags of cotton. 50 bags of cotton. He asked Mr. B, can you please keep these cotton in your godown? He said yes. Of course, bailment now. Okay. While the goods were in the warehouse, that day there was a huge rain and it flooded. Of course, the 50 bags of cotton was destroyed. Now the question is, who will bear the loss? Is it the bailer or the bailee? Yes, you guys are right. It will be bailer's responsibility. Act of God. I have taken reasonable care. I have kept it in a warehouse. Even after that, if it rains, what else I can do? So act of God, something which is not in my hand, after taking reasonable care, even if some damage happens, it will be the responsibility of the bailer. Bailee will not be responsible. If I have taken proper care of the goods, I will not be responsible. Shantilal versus Tara Chanda Madan Gopal. Unit 9, last one of Indian Contract Act. Anoda Persad Roy versus Dwarkanath Gangopadhyay. Now in this case, what happened, people? Of course, as an agent, people, you need to give proper accounts to your principal. What do you mean by proper accounts? Proper accounts means the numbers, journals, ledgers supported by vouchers, deeds, invoices. That's the meaning of supported by proper documents. Meaning you have to give render proper accounts means what? Not just giving some journal entry. You have to give supporting documents also, is what was decided in this case law. Exam point of view, okay, not that important. Done Indian Contract Act. Next we are starting with Sale of Goods Act. Directly we are going to Unit 2. Unit 1, no cases. So priest versus last. What is this, people? Whenever I have made quality or fitness, people, whenever I have told you my usage. So in this case, what happened? A went to a shop and said, I want to buy a flask. Now, why do we buy a flask? Flask is always purchased to keep hot water or cold water. So the person relied upon the judgment of the chemist, meaning the shopkeeper. So I told you my purpose and I relied upon your judgment. You gave a product. He went to home and poured boiling water, people. The water exploded. So people, it is an implied condition of quality or fitness. If it is not serving my purpose, people, I will hold you liable. So quality or fitness will come into picture, and I have to rely upon your judgment. If I have relied upon your judgment, people, you will be liable. Priest versus last. Implied condition, quality or fitness is the main thing. Bombay Burma Trading Corporation Limited versus Aga Mohammed Khalil Shirazi. Same thing, people. Quality or fitness. I have told you my purpose. So in this case, what happened, people? Meaning railway company, people, they placed an order with a furniture company. They said, we want certain wooden logs. We wanted certain wooden logs for using it as railway sleepers. Now, what do you mean by railway sleepers, people? Don't get confused with railway sleepers. Railway sleepers does not mean seats. Railway sleepers means those which are put on track. We'll have iron track. You can see wooden logs put like this. These are called as sleepers. So now there was a company which supplied these sleepers, people, but it was unfit for it. Why? It rained. The wood spoiled. When the purpose was told, railway sleepers, I know it is outdoor. Who will use it indoor? Da? So it was your duty to give it as per that. Again, people, what is it? It will come under specific purpose when it is communicated. Quality or fitness. It has to serve that purpose. Correct? Done. Unit 3, Lee versus Butler. Meaning what, people? Okay, case only. What is this? A told B that I'm selling my goods to you on hire purchase agreement. You have to pay me monthly installments. So this was there in the condition. It is hire purchase, it seems, and you have to pay me money on installments. And remember, you can never terminate the contract in between. Meaning you have to pay. You don't have a choice of going back. The question is, people, A gave goods to B. B further sold this goods to C. The question is this, people, is this a valid sale? Remember, if it is a hire purchase, people, until the last installment is paid, you can never become the owner. So in a hire purchase, sub-sale can never happen. So it will not be considered as a valid sale. But in this case, people, the seller had put one condition. What? It's a hire purchase agreement. It was written. Correct. Valid. But they had put one more condition also, people, that you cannot terminate the contract in between. Remember, hire purchase agreement can be terminated if any installment is not made. So the contract, the court read it as, even though you have named the contract as hire purchase, but the effect was not like that. The conditions was not like that. So they considered this contract not as a hire purchase. They considered it as a conditional sale and not as a hire purchase, even though you have named it, because your terms was not that of a hire purchase, and the sale made by B to C was considered as valid. Exam point of view, no, they won't. Mount DF Limited versus J&J Provisions, Unit 4. What are those, people? Nothing but sub-sale. Is it valid? Yes. A sold goods to B. B said, I don't have money now. I will further sell it to C. Whatever they pay, from that I will pay to you. Now, A sold, ownership was passed. This person also paid money, but this person did not pay the money. The question is, this person's right as unpaid seller, will it come to an end or will it continue? The answer is, people, remember, whenever you have agreed for a sub-sale, whether directly or indirectly, people, your right as an unpaid seller will come to an end. So this will be a valid sale. Mount DF Limited versus J&J Provisions. I hope it is clear. Done. Chapter 4, Unit 1. Nothing but Indian partnership, no much cases here. Santiranjan Das Gupta versus Dasiran Murzamul, KD Kamath and Co versus CIT. Both the cases, the case is on simple thing, whether is partnership there between the parties or not. So the court saw a lot of aspects and decided what is the true test of partnership. So whenever you're writing this case law, the main word provision you will be writing this case law for will be this true test of partnership. What and all will be seen? Of course, people, mutual agency, presence of bank accounts, profit sharing, business being present. A lot of things will be considered, and then only it will be said whether this is a partnership firm or not. Was what was decided in both the case laws. So whenever they're asking you any question on true test of partnership, then please feel free to quote in these two. This will be a superior case law. One is sufficient. So remember and go. More than sufficient. Unit 2, Vishnu Chandra versus Chandrika Prasad. In a partnership deed, there was one clause which said, a deed saying if they wants to dissociate from the partnership business. Meaning what, sir? If at all a person wants to disassociate from the partnership, meaning he wants to leave, he needs to give a notice. Now the question was, the words disassociate from the partnership. Let us imagine, are they referring to if A, B and C, if C wants to go away, he needs to give a notice? Is that what they are trying to tell? Or are they telling if C wants to put an end to the complete partnership firm, complete disassociation, he needs to give a notice? What is that they are trying to tell? Is it they are trying to tell if C gives a notice, he can go, or if C gives a notice, entire partnership firm will be dissolved? What is the intention of that word given in that agreement? The court interpreted it as they meant to say it is one partner going out, that is the intention, and not the entire firm coming to an end. Exam point of view, not important. Makora versus Northern Assurance Company Limited. What happened in this case? There was a person, Companies Act we have started, people. There was a person who has taken insurance on all the company's assets. All the assets of the company. But he has nominated himself as a nominee. So one day it so happened that all the assets of the company, there was a fire breakout. But when they went into the case, it was seen that this person has tried to show that assets belong to him and not to the company. And in this case, it was decided that separate legal entity concept, the assets will belong to the company, the money will also belong to the company only. So the contract was not validly taken. If you remember, people, contract of Uberima Fidus, you cannot hide any detail. Misrepresentations cannot happen. It will be fraud. So the contract was not valid and not binding on the insurance company. Was what this case law, Makaura versus Northern Assurance Company Limited. You will quote this case law for, you will quote it for what? Separate legal entity. Next one, of course, same case law, Salomon versus Salomon also. Whenever a company is formed, what happened in this case law? A person formed a company. A person formed a company. Now, this person is called as Salomon. So, he is also a shareholder in the company. And when a company wanted some money, after some time, company wanted some money. The company went and borrowed the money from banks also. And the company had borrowed money long back from this person also, Salomon also. So, Salomon also had given the company some money. So, the company had to repay loan to both. One is to outsiders, one is to Salomon. But Salomon people called himself as a secured creditor. Meaning what? Whenever repayment happens, the first priority will always be given to a secured creditor and not an unsecured creditor. So one fine day, the company went into liquidation. The company does not have sufficient money. Imagine like this, the company has 5,000 rupees left with it. In that 5,000, they have to give bankers 10,000 and they have to give Salomon another 10,000. But the money left with the company is only 5,000. who should the company give the money to? The bank said, hey Salomon, you and your company are one and the same. It is your responsibility to give the money to the outsiders first and then you take. In this case, it was decided, people, once the company is formed, it has a separate legal entity. It enjoys its own existence. So bank and Salomon both are the same for the company. Both of them are outsiders. And the bank's loan was unsecured. And the Salomon's loan was secured. So Salomon enjoyed the priority. So he took the 5,000 rupees. Again, it is a principle. What is the main fact for? What is the conclusion? When you're writing the provision is for separate legal entity. Important from company law's point of view. Simple, done, done. Next one, Daimler Company Limited versus Continental Rubber Tires. This is a case law for people lifting of corporate wheel. Generally, people separate legal entity means company is different and shareholders are different. But whenever a company form of business is utilized to do something which is, fraudulent, unlawful, in such cases, people, we will lift the corporate wheel and we will say company and the shareholders are one and the same. One such case is, people, Daimler Company Limited versus Continental Tire and Rubber Company. In this case, what happened, people? There were certain citizens in Germany. There were some citizens in Germany. They opened a company. They incorporated a company in UK. This was into manufacturing tires. This company was supplying tires to another company in UK. All of a sudden, this company started saying, we do not want to buy the tires from your company. After having a 5-year contract, they started saying, we don't want your tires after 2 years. So when questioned why, the matter went to court. So they said, sir, we do not want to buy tires from this company because they are our alien enemies. But the company incorporated in UK said, let us imagine company A said, sir, we are not alien enemies. We are also registered in UK. They are also registered in UK. Why are we alien enemies? So company B said, no, sir. They are not alien enemies, but their shareholders are alien enemies. But company A said, sir, we are registered in UK. Separate legal entity, no. They are different. We are different. But company B proved that, people, sir, let us agree. What they said is true. And we will give money to this contractor. We will give mast money. Then, people, the company will start earning more and more profits. That time company will declare dividends. That means indirectly the money is going for German. People, this was happening during the World War time, people, where Germans and UK citizens had declared each other as their alien enemies. So in the court, it was decided that when the corporate wheel is lifted, the company and the shareholders are same. The corporate wheel was lifted. Yes, the company set aside this contract. Done, done. Jaggilal Kamlapat, Commissioner of Income Tax. What are these people? If you guys remember, we had seen one case in our class, Dinsha Manekji Petit. What happened, people? This case, simple, people. One person formed a lot of companies he formed. Imagine, people, now I have money. Let us imagine I have 1 lakh rupees. If I directly invest in Infosys will declare me dividends. Now, whenever Infosys declares dividends, it's an income for me and hence I need to pay tax. Yes. So anyone would do it in the same way. But what did this person do? This also is called a case of Dinsha Manekji Petit. Same case, same facts also. What this person did? This person formed 3 dummy companies, shell companies, no activity at all. So whatever 1 lakh rupees he had, he further divided that money into various companies. Like I gave 40k, 30k to these companies. What will this company do? This company will further invest in various companies like Infosys, Tata, ITC. Now they are all dividend giving stocks. They will give dividend every year. They started giving dividends to these companies. So this company started earning profits. That means they should pay tax as per this country's rules. Now what did this person do in the top? Mastermind. He started taking all the profits that the companies made. He started taking those profits as loan. He started taking it. And he never repaid the loans to these companies because it is his companies only. 100% of shareholding was with him only. He never repaid. By which people, what did he do? He did tax evasion. Neither the companies paid. Neither did he pay. Why will he pay? What he got is loan. Will anyone pay tax on loan? No one will pay, no. So what did he do? He came up with a structure to evade tax. So in this case, it was decided, people, if at all. Now what happened? He never repaid the loan also. For these companies, it became bad debts. So no profit. Then no tax. So people, corporate wheel was lifted and said, this person and these dummy companies are one and the same. Whatever profits was made by this company, this person has to pay tax on it. Case law, Jaggilal Kamlapat versus Commissioner of Income Tax. Done. Yes, sir. Again, one more case law, people. Again, lifting of corporate wheel only. Workmen employed in Associated Rubber Industries Limited versus Associated Rubber Industries Limited. What happened in this case law? See here. There was a company A. There was a company B. So, company A had lot of workers. Now, as per the rules of the land, what did it say? Whenever a company earns good profits, whenever you earn good profit, it is of course because of your workers' hard work. Because of them only you would have earned money. So the rule said, people, whenever you make good profits, it is your duty to give good salaries, good commission to your employees also as bonus. Company A had also done some investments in various companies. I'm just giving you an example of one company. Now, of course, whenever I invest, even they will also give me returns like dividends, interest and all, because of which again my profits are going up. If my profit goes up, I should again give it back to my employees also. So what did company A do? Company A came up with a mastermind. They formed one dummy company called as company C. And whatever investments they made in company A's name, they transferred, they sold all that shares to company C. Now, who is the shareholder in company B? Not company A, company C. Now, all the dividends started going to company C, by which company A's profits started falling compared to previous year. The bonus of the employees also started falling compared to the previous year. Now the question is whether whatever the company did, the company C, is this valid or invalid? In this case, it was decided there is no difference between company A and company C. Company C was just created to evade some statutory obligation that is there in the law. So statutory obligation is nothing but people payment of bonus. To evade that, you created this dummy company, and hence these two people are one and the same. Corporate wheel lifted, people, and hence you are liable to give commission even on the profits earned by company C. Was the case law. Associated Rubber Industries case. Then next one. Merchandise Transport Limited versus British Transport Commission. What are the case law? Simple case law. Company A applied for certain licenses of its vehicles with British Transport Commission, like our RTO office. But there were some irregularities because of which the British Transport Commission cancelled the licenses of these vehicles forever in the name of Company A. Now, Company A, of course, cannot shut down their business. What did they do? They formed a subsidiary company. Because what did BTC say? In your name, you can never apply for licenses again going forward. So what did Company A do? Company A formed another company, subsidiary company, Company B. They applied for a license again in its subsidiary company's name. The British Transport Commission rejected this also and said, a lifting of corporate wheel. When I said you cannot do directly also, you cannot do it indirectly also. You both are same only. Again, people, lifting of corporate will when a subsidiary is used as an agent of the holding company. Lifting of corporate will, even this license was also rejected. Clear? Next one, sir. Gifford Motor Company Limited versus Horn. Again, lifting of corporate will, people. Meaning, if at all you are trying to evade any provision of law or any legal obligation or any contractual obligation, to avoid it or fraud, if you are entering into any or if you are opening a company, it will be considered as invalid. In this case, what happened, people? A company called as Gifford Motor Company, they hired one person as their managing director, and this person was called as Horn. In his appointment letter, it was clearly written that if at all in the future, if you resign or if we remove you for the next 3 years, you are not supposed to do anything which will make our customers come to you. You are not supposed to do anything. After 6 months of him joining, people, some things did not work out between them, and Horn ended up being removed in the company. Now, what did Horn do? Horn knew everything about this company. He started selling spare parts of the company. Gifford Motor Company sent a warning to Horn. Horn, there was a clear restriction for the next 3 years. You are not supposed to do anything which will make our customers come to you. So, selling us spare parts, our customers are coming to you. You are not supposed to do that. Now, what did Horn do? Horn opened one company. Imagine, people, H Limited. He made the shareholders as his wife and his friend were the shareholders. Whatever he tells people, they will listen. That was the agreement. Now, what happened, people? The company, H Limited, started selling the spare parts of Gifford Motor Company. This time, people, Gifford Motor Company's patience was tested. They filed directly a case against H Limited saying, "Hey, Horn, you are only doing something indirectly." Horn said, "Hey, what are you telling? The restriction was with me. You entered into a clause with me that I am not supposed to attract. H Limited is a separate legal entity. You do not have any agreement with them." In the case, it was decided Horn and H Limited are one and the same. This person is trying to do something indirectly. And hence, people, in this case, lifting of corporate will to avoid some contractual obligation to do fraud. Lifting of, see, these cases, cut, copy, paste will come here exam. Story also will repeat. Are you getting? If I am not wrong, people, from this case law series, you will at least get 10 marks, people. At least I am telling you. Bare minimum. Yeah? Okay. Next one. Narendra Kumar Agarwal versus Saroj Malu. Exam point of view, not important. Again, lifting of corporate wheel only, people. If at all you guys have formed any company for doing any business which is unlawful, and to find that out, if we want, we can lift the corporate wheel, was what discussed in this particular case law. Not important from exam point of view, but this is the judgment. Separate legal entity to find out unlawful activities being conducted by the company. Lifting of corporate wheel can be done. Simple, done. Harinagar Sugar Mills Limited versus SS Junjunwala. For your level, this case and all is not required at all. But I mean, they've just put it. But yes, what is this case, people? Remember, it's nothing but in a company, people, there will be two types of shareholders. One is called as majority shareholders. One is called as minority shareholders. Majority means, people, let us imagine Reliance, the promoters, Mukesh Ambani family is majority shareholders. Rest of us, like public, we can be considered as minority shareholders. Minority shareholders. So, in this case, it was decided, people. Remember, generally the company will always follow whatever the majority shareholders say, because they will be holding 75% of it, no doubt. But is it always like that? Whatever majority says, should we always follow that only? Should we completely ignore minority? The answer is no. In Companies Act 2013, earlier and all, yes, that was the case. Whatever majority say, that will only prevail. But in Companies Act 2013, that is not the case. Whatever minority says, even that will also prevail as long as they are right. So even minority shareholders are also given right to speak. This is under Companies Act 2013. For your level, not at all required. Yes. State Trading Corporation of India Limited versus Commercial Tax Officer Visakhapatnam. In this case, what happened? Okay, I'll tell you what is the summary. The summary was, people, the question in this particular case was whether you guys are considering company as a separate legal person. Agreed? Yes, it's a separate legal person. First of all, is company considered as a person? Yes, it's an artificial person. Now my question is, if I am a person, now Sai Kumar, me, I enjoy something called as people fundamental rights as a citizen of India. Now the question is, people, will the fundamental rights, can even a company enjoy? Forget about that. Can even, okay, I am considered as citizen of India. Can a company be considered as citizen of India? You're a person like me. Can you be considered a citizen like me? In this case, it was decided. Remember, citizenship is only for individuals and not for corporates. That's all. And hence, can you enjoy fundamental rights? No. It is only for citizens, not for corporates. So a company cannot be considered a citizen, and hence you cannot enjoy any fundamental rights given in the Constitution of India. Exam point of view, not that important. Spencer and Company Limited versus Commissioner of Wealth Tax. What happened, people, in this? Again, people, same thing. Dinshaw Manekji Petit, same thing. Evasion of tax, lifting of corporate wheel. Nothing else will change. So Spencer and Company Limited versus Commissioner of Wealth Tax. Cut, copy, paste. So whenever they're asking you for evasion of tax, feel free to write this case law. It will be valid. Spencer and Company Limited versus Commissioner of Wealth Tax. Heavy Engineering Mazdoor Union versus State of Bihar. Sir, in this case, what happened, people? Sir, there is a central government, sir. Central government is holding 55% of shares in a company called XYZ Limited. Now, we all know that this is a government company. Yes. Now, my question is, people, the workers of this government company, should we consider them as government employees? Should you consider them as government employees because they are working for government only, no? Central government only, no? Remember, people, even though you are a government company, you will not be considered as government employee. That means what, people? You cannot consider XYZ Limited as government only. When the company is incorporated, it is a separate legal entity. You cannot consider XYZ Limited as government. It's a government company. End of the day, company only. That means what? You cannot consider it as one of the, you cannot consider it as also one of the government. So I cannot consider them as government employees, and hence pension, all those rules will not apply. So in this case, there was a fight and argument that when a shares are held by government in a government company, then that government company will also be considered as government. And hence all the employees will be government employees. And whatever laws applies to government will apply to government company also. Answer is no. It's end of the day company which is held by government. The employees will not become government employees, and all that was what was decided in this case law. Case law, again, principle is for separate legal entity. No matter whether you are the shareholder or government is the shareholder, company is company only. Clear? Separate from its shareholder. Borland's trustee versus Steel Brothers and Company Limited. In this case, what was decided? Again, not required for us, but people, doctrine of constructive notice. In this case, what happened, people? A shareholder had once the articles of association is registered, the shareholders are bound to the company. So in the articles of association, people, there was one rule. What does it say? That if a company, imagine if a person becomes insolvent at any given point of time, if a person becomes insolvent, at what price the shares should be sold will be decided by the company and not by the insolvent. This condition was there in the articles of association. So just like that, people, a person became insolvent also. So on behalf of him, an official liquidator was appointed to come and sell all the shares of this person. All the assets of this person. One of the asset was also shares. So the official liquidator wanted to sell the shares at 150 rupees per share. But the company said, no, nothing doing. You cannot sell it more than 100 rupees per share. So the company said, no, we have clearly written in articles of association, you cannot go beyond what is given in articles. The liquidator is coming and saying that, no, it's my right. When I have a share, it is my right. I will sell it at whatever price I want. You as a company cannot dictate it. In this case, it was decided, people, remember, whenever the articles of associations is registered, the shareholders are bound to the company. The company is bound to the shareholders. Whatever is written in articles of association, you are bound by it. And hence, yes, in this case, you cannot sell for a price higher than 100, which is given in our articles of association. And you are bound by it. That is what was discussed and decided in this case law. Exam point of view, okay, not that important, you can ignore. Ashbury Railway Carriage Company and Iron Company Limited. What is this, people? Doctrine of ultra vires. Simple, I'll tell you in other terms. Imagine, sir, there was a company whose articles of, whose MOA, object clause said we can do any contract which is railway construction, railway contracts, all that we can enter into. The directors of a company entered into a contract to give loan for someone else to build a railway company. So our directors enter into a contract to give loan to build a railway company to someone else. What did we give? We gave a loan. The shareholders came and said, people, whatever you guys entered into a contract to give loan to the railway company is ultra vires. The directors are saying, no, how is that? How is it ultra vires? It cannot be considered as ultra vires. Because, people, what has happened here? How can it be considered as ultra vires, people? Yeah, directors are trying to say that it is not considered as ultra vires transaction. But people, remember, end of the day, we are giving loan for a other company to build a railway company. Giving loan is a finance transaction, which can be done only by people, a banking company. So did the directors, whatever they do, was it valid? Answer is no, people. It was a ultra vires transaction. They went beyond their object clause. And hence it does not bind the company. It is an ultra vires transaction. Understood? Again, Tamte started. Okay, next case, people. Royal British Bank versus Turkey. In this case, what happened, people? The company, in its articles of association, has clearly written the company's directors cannot borrow loan beyond an amount given and agreed in the company's shareholders meeting. Whatever is the maximum limit agreed in the shareholders meeting, whatever is the maximum limit that is agreed by the shareholders in the meeting, the company cannot borrow. What nonsense.
It was audible there. Yeah. So it was clearly given, people, in the articles of association that the company cannot borrow, the directors cannot borrow loan beyond the number that is mentioned in the company's general meeting. Whatever the shareholders have authorized in the general meeting, the directors cannot borrow money beyond that. So where will it be agreed? It will be agreed in the general meeting of the shareholders. But wonder what happened, people? The directors of the company went and borrowed money from a bank called as Royal British Bank. How much did they borrow? They borrowed, let us imagine, 10 lakh rupees, which is repayment of 1 year. After 1 year, people, 1 year is done, the company did not repay the money. The company did not repay the money. Now the question was, people, what did the company say? When the Royal British Bank came for asking the money back, the company said, people, sir, so sorry, we are not liable to pay 10 lakh because the money that we had authorized in our general meeting was only 5 lakh. Why did you guys give our directors beyond 5 lakh? So people, in this case, it was decided, people, that are the outsiders allowed to attend your meetings? No. So how will they be aware of whatever was discussed in your meetings? So people, in this case, it was decided, people, the company will not, the bank, the outsiders will not be liable for whatever they are not aware of, and that is only called as, people, doctrine of indoor management. Outsiders are not allowed to come into this meeting. So how will I know what was agreed in this meeting? So what would be the right way? The right way is, people, to put it in AOA. Say that your directors cannot borrow beyond 5 lakh. Put it there. Yes? Agreed? Yes. So in this case, the bank was able to recover the money under the rule of doctrine of indoor management. Next one, people. Ganesha. I hope you guys are able to hear that background noise. You guys are in the background there, when 500 speakers are playing top 10. I hope you guys are not listening to that. The voice is not. SS Rajkumar versus Perfect Castings Private Limited. In this case, what happened, people? Nothing but a contract was entered into violation of restriction in the articles. When challenged, the outsider argued that they were unaware of the restrictions. What is that? A company's directors entered into a contract with the outsider in violation of its articles of association. So when challenged in the court, they said that as an outsiders, we do not know what is there in the articles. How will we know? Doctrine of constructive notice, people, ignorance of law is not an excuse. If the documents are sitting in the public domain, whether you read it or not, it is always understood that you have read the documents. Principle, people, doctrine of constructive notice. Howard versus Patent Ivory Manufacturing Company Limited. What is this, people? This is a case for exception of doctrine of indoor management. What is this, people? Nothing but in a company shareholders meeting, it was decided that a company cannot, the directors cannot borrow any loan without asking shareholders beyond 5 lakh rupees. Was it given in AOA? No. Was it given in MOA? No. But where was it written? It was nowhere written, but it was decided in the shareholders meeting, for which even the directors are also one of the participants. They also participate. No. Now in this case, what happened, people? When the company wanted money, one of its directors only gave loan. 10 lakh rupees was given by the director to the company. The question is, people, he said that's a doctrine of indoor management. In this case, it was said, people, it does not protect the person who is aware, who is having the knowledge of the irregularity. You know that you are not supposed to borrow more than 5 lakh. You are aware of it. And if you give 10 lakh, people, whether the company will be, liable to pay it or not, you are aware of it. In the previous case, Karkan's rule, it was outsider. Here you are aware. And you are not entitled for the money back. It is only 5 lakh rupees. But remember, I told you in Mohri BB case also, there is something called as doctrine of equity. If company has taken the benefit, people, it is your responsibility to return that. You cannot say, I will take benefit of 10 lakh and I am not liable to repay. That you cannot say. That will always be your right. And it is your liability. Clear? Morris versus Canson. Nothing but, people, this is same. Morris versus Cranston is the same case law for Rubin versus Great Bengal Consolidated. What is that, people? Exception to indoor management. In this case, what happened? One of the person applied for some shares in the company. One of the person applied for some shares in the company. In that company, there was one secretary. This person did a forgery of the signature of their directors. And he issued the share certificate to this person. Later, when the company got to know, they said, no, this transaction is invalid. He is an innocent buyer. Now, the question was whether he will get the shares or not. So, in this case, it was decided, people, always remember, forgery will never give anyone a right. You can file a case on the secretary, that's a different story, but the company will not be liable or responsible for this act. So whether will this be liable? Answer is no, it will not bind the company. Exception to doctrine of indoor management. No matter how innocent you are, company will not be liable for this contract. Is clear? That is Rubin versus Great Bengal Consolidated. Same thing is this also. Which one? Morris versus Cranston. Ignore this. Remember Rubin versus Great Bengal Consolidated. Next one, people. Anand Bihari Lal versus Dinsha and Co. Again, one of the example for people. Your exception of doctrine of indoor management is nothing but suspicion of irregularity. Meaning what, people? Whenever you guys are entering into a contract with a company. In this case, what happened? One person wanted to buy a property from a company. He wanted to buy a property from a company. He went and gave money. He entered into a contract. He signed everything. Contract, everything was made on behalf of the company by a person. And who is this person? This person is an accountant. Now, people, it is your duty to check people whether with whomsoever you guys are entering into a contract, it is your duty to check whether that person has a right to enter into a contract on behalf of a company or not. You cannot say doctrine of indoor management for everything. In this case, the accountant of the company sold the property to an outsider. Can it bind the company? Answer is no, exception to doctrine of indoor management. Case law, people, Anand Bihari Lal versus Dinsha and Co. And the last case, people, is Horton and Co. versus Northern Law and Wills Limited. Nothing but, people, case law is similar to whatever is seen in Anand Bihari Lal. Notice of irregularity. Meaning, people, when you know that something is not right and you have not made your enough research, in such case, companies will not be held liable. That is these cases, and luckily we are done. In the background, I don't know, they are going to kill me with the sound, I think so. I don't know why all this, but yes. Okay. Hopefully, yes, the same God, or the God, whatever we believe in, hopefully gives us the marks that we guys expect and anticipate. And I hope this session made some sense to you. And I'm screaming here because of the background music. But do let me know your comments. I'll be the most happiest person to know how it helped you. And wish you guys the best in tomorrow, day after tomorrow. Let us do your RTPs and MTPs. And the last day will be for the practicing of your writing answers. So thank you so much, people. I hope it was a very good quick revision of all the cases that is there in your ACCA syllabus. Thank you. See you all. Bye-bye.
Hello guys. Hope you are able to see. I hope everything is working fine. If you guys have any doubts, I thought, yes, why not directly go live? And yes, if you guys have any doubts, we can discuss that as well. And yep, let us, without any delay, let us start with your RTPs. I hope you guys have done with your last 3 days schedule, whatever we are done. And that part is sorted is what I believe. But if you guys have any doubts, you can please let me know and I'll try to answer that. So to start that, I got the last 5 RTPs. Yep. More or less, in certain places I'll try to tell you that these are the important topics. Try to remember them because they have repeatedly asked them. Based on that only I've prepared the most important topics as well. So make sure you guys watch that most important topics part. Do not skip that at any cost. It is very, very important because on that we see a lot of questions being framed. Yes, so do not skip that part. And I hope I'm audible to all of you. So let's start. So wherever possible, you guys also try to answer and you will understand where you guys stand. Yeah. Okay, we'll start. Mr. Parth applied for a job as principal of a school. The school management decided to appoint him. One member of the school management committee privately informed Mr. Parth that he was appointed, but official communication was not given by the school. Later, the management of the school decided to appoint someone else as a principal. Mr. Parth filed a suit against the school for cancellation of his appointment and claimed damages for loss of salary. State with reasons. Will Mr. Parth be successful in suit filed against a school under Indian Contract Act? So people, it is clear. It is rules of acceptance. The acceptance here was not formal. It was informal. Point 1. Point 2, people. Acceptance should always be given by the person that is promisee. He should give the acceptance or any other person authorized by him. A random person cannot give an acceptance, right? If I have made an offer to you, you have to give an acceptance, or if it's a general, then anyone can give. But in school, it's not like an attendant, a clerk, a student, or a parent sitting there. They cannot give an acceptance, right? It has to come from a formal person. It has to be by a promisee, or it has to be by a person, any other person authorized by him. So on that ground, I can tell people this is not a valid contract and you will not get any right in this particular suit. So my answer will be whether Mr. Parth be successful? Absolutely no. He will be unsuccessful. That will be my conclusion. I will write in conclusion, Parth will not be successful, referring to my provision. Clear? Rules of acceptance. Sarthak is employed as a cashier on a monthly salary of 50,000 by ABC Bank for a period of 3 years. Mohit gave surety for Sarthak's good conduct. After 9 months, the financial position of the bank deteriorates. Then Sarthak agrees to accept a lower salary of 40,000. So earlier the guarantee was given for 50,000 salary. Now it has become 40,000. Okay, per month from the bank. 2 months later, it was found that Sarthak had misappropriated cash from time of his appointment. What is the liability of Mohit taking into account the provisions of Indian Contract Act? Hi Nandu, hi Nitin, hi Sai Charan. Yeah, hello. So in this case, what happens, sir? If you guys remember, people, the question is coming from your indemnity and guarantee. In guarantee contracts, whenever there is any change in the contract between, we would have seen it like this. If at all there is any change between, imagine, principal debtor and the creditor. If at all there is any change between them, and if it is not informed to the surety, to the guarantee, if any material change happens, people, then the surety will be discharged from the contract. So in this case, there has been a material variance, people. There has been a change in the contract which is not yet intimated to the surety. The guarantee is not yet intimated, and that will be my provision. So my conclusion, what will be my conclusion? My conclusion will be, people, in this case, what they're asking you, what will be the liability of Mohit? Mohit is who? The surety. The liability of Mohit has come to an end because of variance in the contract without the consent of the surety. That will be my conclusion. I hope this is clear. Hello, David. Yeah, Rahul was, I hope that is clear. Are you getting how I'm phrasing my answer? Are you getting? My first part will always be provision. My last part will always be conclusion. Opening statement should be law always. Are you getting my point? Yes? Hello, Navya. Rahul was a DJ at a 5-star hotel. DJ Macha. As per the contract, he is supposed to perform every weekend. Okay. That is twice a week. Rahul will be paid 2,500 rupees per day. However, after a month, Rahul willfully absents himself from the performance. Taking into account the provision of Indian Contract Act, you have to answer these three following. People, whenever there is one question with three answers, and if the question is belonging to a same provision, have one provision and write a conclusion like this: 1, 2, 3. So my provision is same here. What is this? Breach of contract. Does the hotel have the right to end the contract? Does the hotel have the right to end the contract? Does the hotel have a right? Answer is yes. Because if you failure to perform the contract, this person did not show up. Can I end? Answer is yes. If the hotel sends out a mail to Rahul that they are interested to continue the contract and Rahul accepts, can the hotel resign the contract after a month on this ground subsequently? People, always remember, breach of contract, failure to perform the contract. I have a right to cancel the contract or continue the contract either by express words or by conduct. I can continue. But once I continue, people, later on, I cannot cancel the contract for the same grounds. So here, once I continue, I cannot cancel the contract. I cannot go back to the contract. Correct? Sir, provide the answer in writing. Rakesh, tomorrow, the last day will be only practicing answers. We will be practicing on how to write. Now today I'll have to do what? We are thinking of doing 5 MTPs. In one MTP, 23 questions are there. So put together will be what? 120 questions. So today I'll not be able to write and practice, but tomorrow's session is for that. We will be practicing and writing. Is this clear? Sir, we are scared about law only. Thank you for your efforts. I know that the law has been scaring all of you guys. That is why every day I've given you a schedule so that you guys will learn the subject with me and you will also be able to finish the subject with me. Yeah. See, consistency, persistence, people, will make you guys flourish. The third thing where I am trying to come, these two are with you. Consistency and persistence is with you. What you do the result will give you. The third thing is, people, the lack of aim. So you want to do, but you don't know what to do. And that is the reason every day I'm trying to come and tell you, do this, it will help. Do this, it will help. So if you guys have been looking at whatever the videos I've been uploading, you just see your past papers, you see past RTPs, you see now past MTPs. The topics that is repeating, the common topics are coming. So the chances of these questions coming again in your exam is always there, 100%. That's why I'm saying no more questions and go. Like now, just sit back. I'm reading the question. You try to predict your answer sitting there. And I'll tell you whether it is right or wrong. Correct? In which of the case, termination of contract or continuance of contract, can the hotel claim damages? So remember, people, either the hotel, whenever there is a breach of contract, what are the two remedies you have? You can cancel the contract immediately, or you can continue the contract. In either case, people, you have a right to claim compensation. So in this case, the company, the hotel has a right to claim compensation in both the cases. Clear? Clear? Bhagya sir, abki bar paper tough aayega kya? No, Bhagya, it will not be tough and all. Why don't we prepare to the toughest paper and then paper turns out to be the most easiest one? Correct? Examine whether the following constitute a contract of bailment or not. So what is bailment, people? Temporary transfer of possession of goods from one person to another person. Once the objective is achieved, the goods will be transferred back or disposed of according to the instructions. So Vikas parks his car at a parking lot, locks it and keeps the keys with himself. People, remember, this is not transfer of possession. It is just a transfer of custody. The car is still under your control and hence this is not considered as bailment. It is just a transfer of custody. Next one, seizure of goods by customs authorities. Of course, they have seized it. The control is with them now. Yes, this will amount to bailment. Clear? Sir, May 25 maths was tough now. Nothing like that, people. We'll now when we are doing so much, then why paper will be difficult? Let us make sure we prepare to the toughest extent, no? Yeah. Mr. Sanjay Kothari was a big businessman having two sons, it seems, and one married daughter. Okay. He decided to gift his house to his daughter. Okay. For this purpose, he called his lawyer at his house and made a written document. See, when you're reading the question only, you should know there is a son, there is daughter, there is a house, there is a written document. Now, I'll not even read the next 5 lines. What will be the question be on? Question will be on exceptions to quid pro quo, natural love and affection. Yes. Written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going for registration of the document, they met an accident and both died. Later, the daughter found the document and claimed the house. Explain whether she can get the house as gift under the Indian Contract Act. Answer is no. Because people, I'll tell you 3 reasons why this is not gift, but why it is considered as a love and affection. Because people, when the parties stand in a near relationship, father and daughter, when the document is written, people, it should be registered, people, and only then it can come under exceptions to quid pro quo. A contract without consideration will be valid if at all it is entered between a near relationship, and if it is for what is that? Natural love and affection, and people, the document has to be written and registered. Here the document is not yet registered, and hence the daughter cannot claim the house based on this particular document. Is this clear? Okay. Mr. Ayush, the employer, induced his employee Mr. Bobby to sell his 1-room flat to him. See, employer, employee. He induced. See, what is the question on? Undue influence. Correct? At less than the market value to secure promotion. Mr. Bobby sold the flat to Mr. Ayush. Later on, Mr. Bobby changed his mind and decided to sue Mr. Ayush. Examine the validity under Indian Contract Act. Of course, people, undue influence, and hence the contract is voidable. Simple. Mr. Suraj promises Mr. Manoj to paint a family picture for 20,000 and assures to complete his assignment by 15th March 2023. Unfortunately, Mr. Suraj died in a road accident on 1st March 2023 and his assignment remains undone. Can Mr. Manoj bind the legal representative of Mr. Suraj? Who can perform the contract? Who can perform? Promiser himself. When the promiser himself has to perform the contract, whenever the contract involves any special skill, talent, confidence, in such case, only the promiser can perform and legal representative cannot perform. In this case, drawing, painting involves a skill and talent, and hence legal representative will not be liable, and this contract is a void contract because of impossibility of performance, and hence whatever benefit is taken should be returned. So if 20,000 has been taken, you have to return it. Okay. Suppose Mr. Suraj has promised to deliver some photographs to Mr. Manoj, meaning I have taken some photos, it seems. I have said that I will sell that to you. Now people, whether I am there or not, the photographs at my home, I can sell it, right? That does not require any special skill or talent, because it is already taken. It's a photograph, it is already taken. So that, yes, the legal representative will be liable to give it to Mr. Manoj. Yes, you will be liable. Yes, sir. Okay, next one. Rahul, I'll tell you, I think we have such questions also on subsidiary company. We'll take it up when it comes. Prakash reaches a sweet shop and asks for 1 kg of burfi if the sweets are fresh. Seller replies, sir, my all sweets are fresh and of good quality. Prakash agrees to buy on the condition that first he tastes one piece of barfi to check the quality. The seller gives him one piece to taste. Prakash, on finding the quality is good, asks the seller to pack. On reaching the house, Prakash finds that barfi is stale, not fresh, while the piece tasted was fresh. Now Prakash wants to avoid the contract and return the barfi to the seller. State with reasons whether Prakash can avoid the contract. Yes, people, whenever the goods are sold in sample, I gave you one piece of barfi. The bulk has to correspond to the sample. The sweet I tasted in the shop was fresh, but the bulk was stale. It was rotten. So the bulk did not correspond to the sample. See, provision, I'm not telling it like a story. I'm not telling it morally, because of the story I feel this is how I need to write. That's where people go wrong. You should not write the law because you feel so. With provision, you have to support the answer. Goods corresponding to sample did not match with the bulk. On that ground, yes, I can. Will your answer be different if Prakash does not taste the sweets? What if sample was not given at all? My answer will not change because he has claimed that all my sweets are fresh and of good quality. This is called as what? Sale of goods by description, and description is not met if sample is not there. So in that case also my answer will not change. You are liable. I can get my money back. Simple. Okay. Akansh purchased a television set from Arvind, the owner of Gada Electronics, on the condition that first 3 days he check its quality, and if satisfied he will pay for that, otherwise he will return the television set. On the second day, the television set was spoiled due to an earthquake. Arvind demands the price of a television from Akansh, whether Akansh is liable to pay the price. People, sale of goods under sale or return basis. I have 3 days time. In the 3 days, if I have taken proper care of the goods, then my liability as a bailee will come to an end. So in this case, if any unforeseen event happens, earthquake, anything, which is not in my control, so as a buyer, I am not liable because I have 3 days time. The ownership has not yet passed. The ownership, when will it pass? Whenever I've given that consent, or if I keep the goods beyond the return period, or if I do something equivalent to an acceptance. I have not done any of these three, and hence the ownership has not yet passed. So the person, the seller himself is liable. I hope this is clear. They online no. I hope it is clear. Mr. Arun contracted to sell his Swift car to Mr. Nikhil. Both missed to discuss the price of the said Swift car. Later, Mr. Arun refused to sell his Swift car to Mr. Nikhil on the ground that agreement was void, being uncertain about the price. Does Mr. Nikhil have any right against Mr. Arun under Sale of Goods Act? See, if the question is asked under Indian Contract Act, the answer is different. Yes, it will be vague because you have to decide the consideration. But Sale of Goods Act, we clearly have a section 9, that is ascertainment of a price. So people, always remember people, in ascertainment of a price, if the price is not agreed, on that ground, you cannot call the contract as void. You have to pay what is reasonable. So if the buyer pays what is reasonable, then the contract will be valid. This is clear? All of you? Okay, done. Next one. Mr. Shankar sold 1000 kgs wheat to Mr. Ganesh on credit of 3 months. Wheat was to be delivered after 10 days of contract. After 5 days of contract, see, this was there in MTP. At least 2 times it is already given in MTP. Again coming in RTP. Yeah, after 5 days of contract, a friend of Mr. Shankar secretly informed him that Mr. Ganesh may default in payment. On the information of friend, Mr. Shankar applied the right to lien and withheld the delivery. With referring to the provision of Sale of Goods Act, state whether Mr. Shankar was right in his decision. What would be your answer if Mr. Ganesh became insolvent within 5 days of contract? People, right to lien can be exercised when the goods are not sold on credit, or if sold on credit but the credit period is over, or when the buyer becomes insolvent. In this case, the goods are sold on credit of 10 days. but this person is cancelling it in 5th day only. Credit period is not yet over. So people, I do not have a right to lien because he has not yet become an insolvent. You are thinking he may default. It is not yet certain. So the seller here cannot exercise the right to lien because the credit period is not yet over. In the second case, what if he becomes an insolvent? Yes, it gives me a valid right. That time I can cancel the contract. I can. As an unpaid seller, I have a right to exercise lien. Done. Moni and Tony were partners in the firm, Measures Moto and Company. They admitted Sony as a partner in the firm and he is actively engaged in day-to-day activities of the firm. There's a tradition in the firm that all active partners will get a monthly remuneration of 20,000, but no express agreement was there. After admission of Sony in the firm, Moni and Tony continued getting salary from the firm, but no salary was given to Sony from the firm. Sony claimed remuneration. You guys decide whether Sony will get it or not. Your answer should just come like this here. What? Can a partnership firm pay remuneration to the partners? Is it possible? The answer is yes. If your partnership agreement provides. Sorry, in this case, it does not provide. If it is customary in the partnership to pay the remuneration. In our case, it is customary because these two partners have been receiving the remuneration for a very long time. So it has become a custom. On that ground, Sony will also be eligible to claim remuneration. Is this clear? Pakka, 100% done. Mr. Ram and Mr. Rahim are working as teachers in Ishwar Chand Vidyasagar Higher Secondary School, Ababa, and also very good friends. They jointly purchased a flat which was given on rent to Mr. John. It was decided between landlords and tenant that the rent would be 10,000 per month inclusive of electricity bill. It means the bill will be paid by landlords. The landlord by mistake did not pay the electricity bill for the month of 2021. Due to this, the electricity department cut the connection. Mr. John has to pay the electricity bill of 2,800 and 200 as penalty to resume the connection. Mr. John claimed 3,000 from Mr. Ram, but Mr. Ram replied that he is liable only for 1,500. Mr. John said that Mr. Ram and Mr. Rahim are partners, therefore he can claim the full amount from any of the partners. Can he claim, people? If at all it is a partnership that is there between these two people, then you can claim a complete, money from one partner. One person. In this case, answer is no, people. We know for a fact, always remember the chances of question coming between partnership and co-ownership is always high. As a student, if I were a student, I will never skip a topic of co-ownership. So in this case, I will say, no, the person cannot recover the entire 3,000 from one person because it is not a partnership. So it is a co-ownership. So this person will be liable only for 1,500. The other 1,500 should be recovered from the other part of the ownership. And it is not partnership. Is this clear, all of you? Pakka, done. Next one. X and Y were partners in a firm. The firm was dissolved on 12th June. But no public notice was given. Thereafter, X purchased some goods in the firm's name from Z. Z was ignorant of the fact of dissolution of firm. X became insolvent and Z filed a suit against Y for recovery of his amount. People, the partnership's liability will continue until a public notice is given about the dissolution. In this case, the public notice is not given, so the partner's liability will continue until the date of public notice about the dissolution. So partners liable, yes, liable. A, B and C are partners of partnership firm carrying on the business of construction of apartments. B, he who himself was a wholesale dealer of iron bars, was entrusted with the work of selection of iron bars after examining its quality. As a wholesaler, B is well aware of the market condition. Current market price of iron bar for construction is 350 per kg. B already had 1000 kgs of iron bar in stock, which he had purchased before price hike in the market for 200 per kg. He supplied the iron bars to the firm without the firm realizing the purchase cost. is B liable to pay the firm the extra money he made, or he doesn't have to inform the firm as it is his own business and he has not taken any amount more than the current prevailing market price? What is the condition, people? Remember, a partner can never make secret profit. First one. Second one, a partner, if he makes any profit using the firm's connection, using the firm's name, using the firm's network, the partner has to refund that money to the partnership. So here, even though you have not made fraud, but you cannot make a secret profit. Either take the consent and do. If not, people, you are accountable to give that profit made to the partnership. Here, yes, you need to return the profits to the partnership firm, because a partner cannot make a secret profit. Clear? Okay. A and B were friends. Now they have plans of setting up a supermarket in their locality. They are confused as to whether to register as a traditional partnership or LLP. Give the difference between LLP and partnership. Basically, they are asking you the advantages of LLP. Okay, Mr. Dhruv was appointed as an employee of Sun Moon Timber Private Limited on the condition that if he were to leave his employment, he will not solicit the customers of the company. After some time, he was fired from the company. He set up his own business under proprietorship and undercut Sun Moon Timber Private Limited. Can anyone tell me which case law it is? Just by looking at it. The company hired one managing director. In that agreement, there was a condition that people that, when you leave the company, you are not supposed to solicit our customers. Can you tell me which case law it is? Which one? Yes, most of you are correct. They're asking you the case law of what, people? The case law of, people, Clifford Motor Company versus Horn. So whether Horn, whatever the activity he did, is it valid? Absolutely no, people. It is invalid. Fraudulent. Lifting of corporate wheel. So the company and Horn are not different. They are one and the same. That is a case law. Correct? Okay, AK Private Limited has borrowed 36 crore from BK Finance Limited. However, as per MOA, AK Private Limited, the maximum borrowing power of company is 30 crore. Examine whether AK Private Limited is liable to pay this debt. State the remedy, if any, available to BK Finance Limited. So people, in my MOA, it is clearly written I cannot borrow beyond 30 crore. So what is the maximum I'll be liable to? I'll be liable to is 30 crore only, not beyond that. So what is the alternative I have? I can file a case on the directors because it is their fault. Why did they go beyond that? So I can hold the directors liable. And not only that, imagine if the directors are going beyond MOA. What I can do? In your remedies for breach of contract, you would have seen one right you have. The right is for people to get injunction order. Order of injunction, meaning stop the company from going against their MOA. You can get an injunction order. You can stop the directors from doing whatever they're doing. So these are the two remedies. File a complaint against the director, make them personally liable, and you can file an order of injunction. Done. Mike LLC incorporated in Singapore, having an office in Pune, India. Analyze whether Mike LLC would be called a foreign company. Yes, people, a company which is registered outside India, has a place of business in India, conducts a business activity in India, will be considered as foreign company. Negotiable. Sachin brought 1000 kgs of rice from Saurabh for 1,50,000 on 3 months credit. Yes, Rahul, correct. For this purpose, Sachin issued a promissory note to Saurabh on the same date payable after 3 months. On the date of maturity, the promissory note was dishonored. Saurabh filed suit for the recovery of the amount plus fees of advocate paid by him for defending the suit. Referring to the provision of Negotiable Instrument Act, what amount could be recovered from Saurabh? People, I can recover the promissory note money, plus I can recover the advocate fees, plus I can also recover 18% per annum as interest for delay in repaying this money. So these are the amounts that I can recover from the person. Is this clear? I hope all of you are understanding the next one. A purchased a watch from B. Okay. He issued a promissory note to B which was payable on demand, but no specific place for payment was mentioned on it. So where to pay, it is not mentioned. On maturity, B did not present the promissory note for payment. As the promissory note was not duly presented for payment, whether A would be discharged from liability under the provision of Negotiable Instrument Act. Answer is yes, people. When is presentment not required? Whenever the place is not mentioned on the promissory note, I am discharged from presentment, people, and hence I need not have to present. And without presentment itself, people, I can recover my money. Done. Yes, that is my one RTP. Done. Let us quickly do the second one. Explain the type of contract in the following agreements. Okay. Rahul contracts with Banu for the supply of 10 tons of sugar, but before the supply is effected, the factory catches fire and everything is destroyed. What type of contract? What happens to the agreement, people? Void contract. Impossibility of performance. Subsequent impossibility. Contract comes to an end. A coolie in uniform picks up the luggage of Rohan out of the railway station without being asked by Rohan, and Rohan allows him to do so. Implied contract based upon the conduct of the parties. Valid contract. Obligation of finder of lost goods to return to the true owner. Valid contract, people. As per quasi contracts, it's a valid contract. Finder of lost goods. Hello. Next one. Amit, a minor, was studying in a college. On 1st July 2023, he took a loan of 1 lakh from Bhavesh for payment of his college fees. Any money taken by a minor for necessity, his estate will be personally liable. Provision is that. And to purchase books and agree to repay by 31st December. Amit possesses assets worth 9 lakh. My assets are liable. I have 9 lakh. On the due date, Amit fails to pay back the loan to Bhavesh. Bhavesh now wants to recover the loan from Amit out of his assets. Possible? Yes, possible. No doubt, absolutely fine. Mr. Sham, aged 58 years, was employed in a government department. He was going to retire after 2 years. Mr. Dev made a proposal to Mr. Sham to apply for voluntary retirement from his post so that Mr. Dev can be appointed in his place. So he asked the government employee to leave his office and go so that I can be appointed. Mr. Dev offered a sum of 10 lakh as consideration to Mr. Sham to do this retirement. Mr. Sham refused at first instance, but when he evaluated the amount offered as consideration is just double of his cumulative remuneration to be received during the tenure, whether the above agreement is valid. So what happened, people? I have taken money to forcefully retire. Is this contract valid, people? Of course, no. Consideration opposed to public policy. Trafficking of public offices and titles. In that you will see. You cannot sell your public office, meaning you cannot sell your post. You cannot sell your job. If any such contract is made, such agreement will be considered as void. It's a void agreement. Clear? Unlawful to public policy. What will be rights with promisor in the following cases under Indian Contract Act? What will be the rights with the promisor? Sunil promised to bring back Jatin to life again. Possible, Ada. It's a void agreement. You will not succeed. Aman, impossibility of performance. Aman agreed to sell 50 kgs of apples to Raman. The loaded truck left for delivery on 15th March, but due to riots in between reached Raman on 19th March, due to which the apples were rotten. People, whenever there is a breach of contract and if the deterioration during transit, so I am discharged, people, I can hold you liable. The agreement is void. An artist promised to paint on the fixed date for a fixed amount of remuneration, but met with an accident and lost his both hands. In this case, people, I'm clearly saying, people, it's a painting, people. So I'm assuming it's a normal paint and it's not a wall painting. So it's a skill. It's a void contract. So contract will come to an end. A void contract. Abhishek entered into a contract of import of toys from China, but due to disturbance in the relation of both the countries, the import from China were banned. People, void contract due to subsequent change in law. It's a void contract. So contract will come to an end. Seema was running a boutique in New Delhi. She has to deliver some clothes to her friend Kiran, who was putting up an exhibition in Mumbai. Seema delivered the sewing machine and some cloth to a railway company to be delivered at a place where the exhibition was to be held. So they have put it in a railway. Seema expected to earn an exceptional profit from the sales made at this exhibition. However, she did not bring this fact to the notice of the railway authorities, meaning she has just given the sewing machine to railway and she has not said why she is giving. The goods were delivered to the place after the conclusion of the exhibition. The railway authorities did a delay. The goods reached the exhibition later than what was expected. On account of such breach of contract, Seema wanted to sue railway authorities. Can she sue? Answer is yes. But people, not for the profits she has lost, she can sue it for ordinary damages because the special circumstance was not communicated. Hadley versus Baxendale. So whatever is ordinary, directly related, only for that you will be liable and not for what is indirect. Explain any 5 circumstances. Okay. Suraj guarantees Vikas for the transactions to be done between Vikas and Nikhil during the month of March. Vikas supplied goods of 30,000 on 1st March and 20,000 on 3rd of March to Nikhil. On 5th March, Suraj passed away. On 10th March, being ignorant of the death of Suraj, Vikas further supplied 40,000. On default in payment, Nikhil on due date, Vikas sued legal heirs of Suraj for recovery of 19,000. Describe whether legal heirs of Suraj are liable to pay 90,000. People, this is nothing but people, a contract of continuing guarantee. The continuing guarantee will come to an end after the death of a surety. After that day, whatever are the contracts entered, the guarantee will not be liable. So does the legal heirs also will not be liable. So in this case, 40,000 happened after the death. So the liability of the surety will be only to the transactions that took place before the death. That will be people 30,000 and 20,000. So the legal representatives will be liable to the 20,000 and 30,000 and not the 40,000. However, also remember the legal representatives will be liable only to the extent of assets inherited from their ancestors. So what is assets inherited? I have inherited only 45,000 worth. Excuse me. So I'll not be liable for 50,000. My liability will be restricted for 45,000. Mr. Stephen owns a chicken farm near Gurugram where he breeds them and sells eggs and live chicken to retail shops. Mr. Fleming also owns a similar farm near Gurugram doing the same business. Mr. Fleming had to go back to his native place in Australia for 1 year. Native place in Australia, rich fellow. He needed money for travel, so he had to pledge his farm to Mr. Stephen for 1 year and received a deposit of 25 lakh and went away. At that point of time, the stock of live birds was 1 lakh birds and eggs were 10,000. The condition was that when Fleming returns, he will repay the deposit and take possession of his farm with live birds and eggs. This is nothing but people pledge. Also remember, pledge includes bailment. Correct? What do you mean by pledge? Pledge is nothing but bailment of goods for security. It's called as pledge. Agreed? So in this case, what I am telling, I am giving 1 lakh, what is that? Birds. Birds. Okay, 1 lakh birds I am giving and I am giving 10,000 eggs. With the condition that after 1 year I'll come back, I'll give back your money. You have to give back my, what is that? Birds and eggs. Okay. After 1 year, Fleming came back and returned the deposit. So he gave back the 25 lakh. At that time, there were 1,09,000 birds. When I gave it was 1 lakh. Now it is 1,09,000. You should know by now, people, in bailment, any accretion, surplus or profits that are caused of the product that is given by the bailor to bailee, the bailee has to return the accretion, surplus or profits that is caused. So I have to give back this people. I don't have a choice. So I have to give back 1,09,000 also. Along with that, even whatever the eggs, I have to give back everything. Simple, done. What this question now? AB Cloth House, a firm dealing with the wholesale and retail buying and selling of the various kinds of cloths, customized as per the requirement of the customers. They dealt with silk, organdy, okay, cotton, khadi, chiffon, and many other different varieties of cloth. Miss Rima, a customer, came to the shop and asked for a specific type of cloth suitable for making a suit for her daughter's birthday. See, she came to the shop and asked for a specific type of cloth suitable for making a suit. People, this is nothing but implied condition as to quality or fitness. Meaning, when I've asked, it should serve my purpose and I should have relied upon your decision. Specifically mentioned that she required a cotton silk cloth which is best suited for the purpose. The shop owner agreed and arranged the cloth piece cut into as per the buyer's requirement. When Rima went to the tailor to get the suit stitched, she found that the seller has supplied her cotton organdy material. The cloth was not suitable for the said purpose. It was heavily starched and not suitable for making the suit at all. The tailor asked Rima to return the cotton organdy cloth as it would have not met the requirement. The shop owner refused to return. People, KVA tempter, as I told you people, I can get back my money because it did not fit my purpose. Quality or fitness, I did not serve my purpose for what I have asked for. Hence, I can get back my money. Samuel purchased a television set from Arun, the owner of Gada Electronics, on condition that people same thing. Again, it is repeating. I'll not again go through. Suraj sold his car to Sohan for 1,75,000. After inspection and satisfaction, Sohan paid 75,000 and took possession of car and promised to pay remaining amount within a month. Later on, Sohan refuses to give the remaining amount on the ground that the car was not in good condition. Advised Suraj as to the remedy available him against Sohan under the Sale of Goods Act. After inspection satisfaction, Sohan paid 75,000 and took possession of the car and promised to pay the remaining amount within a month. Later on, Sohan refuses to give the remaining amount on the grounds that the car was not in good condition. Advised Suraj as to what remedies available to him against Sohan under the Sale of Goods Act. People, unpaid seller people, I have a right to recover for the suit of the price. That is, I can recover 1 lakh. If he doesn't pay, I can recover the legal cost. I can also recover it with interest. That's all. Remedies available against the buyer. Akash purchased 100 kgs of wheat from Bhaskar at 80 rupees per kg. Bhaskar says that wheat is in his warehouse in the custody of Kishore, the warehouse keeper. Kishore confirmed to Akash that he can take the delivery of wheat from him, and till then he is holding the wheat on Akash's behalf. Before Akash picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now Akash wants his price on the contention that no delivery has taken place. People, nothing but the delivery can be of how many types? Deliveries of how many types? There are 3 types of delivery. One is what? What? Delivery, what are the different types of delivery? Delivery, symbolic delivery, constructive delivery. The question is, people, constructive delivery. So, acknowledgement. So, one person said, I am holding the goods on your behalf. So, it's a constructive delivery. The delivery has happened. You cannot recover the price. Sahil, Amit and Kunal were partners in a firm. The firm is a dealer in office furniture. They have regular dealings with Measures AB and Co. Okay. For the supply of furniture for their business. On 30th June 2023, one of the partners, Mr. Kunal, died in a road accident. The firm ordered Measures AB and Co. to supply the furniture for their business on 25th May 2023. So died after the contract was made. Now Sahil and Amit continue the business in the firm's name after the Kunal's death. The firm did not give any notice about Kunal's death to the company or the person dealing with the firm. Measures AB and Co. delivered the furniture to the firm on 25th July. The fact about the Kunal's death was known to them at the time of delivery of goods. Afterwards, the firm became insolvent and failed to pay the price of furniture to Measures AB and Co. Now, Measures AB and Co. has filed a case against the firm for recovery of the price of furniture. With reference to the provision of Indian Partnership Act, explain whether Kunal's private estate is also liable for the price of furniture purchased by the firm. People, after the death, people, whatever are the contracts, I will not be liable. So after the death of the partner, any contracts entered by the partnership firm, the partner or partner's estate will not be liable. Is clear, all of you? Done. State whether the following are partnerships under the Indian Partnership Act or not. A and B buy commodity X and agree to sell the commodity with sharing the profits equally. People, there are two people. Buying and selling, business is happening. Sharing of profits is happening. Hence, I will call it as partnership. Two firms, each having 12 partners, combined by an agreement into one firm. So, people are coming and they are coming it by an agreement. So, I will call it as a partnership firm. A and B, co-owners, agree to conduct the business in common for profit. A and B, co-owners, but they are agreeing to conduct the business. Generally, why do we say co-ownership is not partnership? Because there will be no business. Here that link, they will do business, it seems. So it is a partnership. Don't write it off as co-ownership alone. Some individuals form an association to which each individual contributes 5,000 annually. The objective is to produce clothes and distribute clothes free. No business, no partnership. A and B co-owners share between themselves the rent derived from a piece of land. No business here. And hence it is just a co-ownership and not partnership. Direct. Okay. A, B and C has decided to set up a new club with name ABC. Basically charitable. So Section 8 company. They plan to do charitable work. Okay. The company obtained the status of Section 8. Okay. However, on 30th September, it was observed that ABC club was violating the objects of the section clause. What powers does CG have? CG has a power to take away, revoke your license, wind up or amalgamate with any other Section 8 company. All that are the rights available to CG. HP Polytech Limited has a paid up capital divided into 6 lakh equity shares of 100 each. 2 lakh equity shares the company are held by central government and 1 lakh 20 are held by government of Maharashtra, that is state government. So 2 lakh plus 1 lakh 20, that is 3 lakh 20. Out of 6 lakh, 3.2 lakh is held by government. Hence it is a government company for sure. No Limit Private Company is incorporated as unlimited company having share capital of 10 lakh. Unlimited company. One of its creditors, Mr. Samuel, filed a suit against a shareholder, Mr. Innocent, for recovery of his debt against No Limit Private Limited. Mr. Innocent has given his plea in the court that he is not liable as he is just a shareholder. Always remember, people, in unlimited company, the creditor cannot directly go and file a case on the shareholder. The creditor has to always file a case against the company first. The company will recover the money and the company will give it to the creditor. And when will the shareholder be liable? The shareholder will be unlimitedly liable only when the company is not in a position to repay the debt. When will you know that? When the company gets into winding up, insolvency, only then I will be unlimitedly liable. So in this case, you cannot directly go and file a case against the shareholder. You have to file a case against the company. Liquidator will be appointed. The liquidator will recover the money from the shareholder and it will be given to the creditor. That's the right way to do it. I hope this is clear. Clear? Hello? Done. Next one. Manoj purchased some goods from Sagar. He issued a check to Sagar for the sale price on 14 June. Sagar presented the check in his bank and his bank informed him on 19 June that the check was returned unpaid due to insufficiency of funds. Sagar sued against Manoj under section 138. State with reasons whether his suit is maintainable. Answer is yes, people. Any legally enforceable debt. If you file a case within 3 months, then yes, people, you can recover the money, because beyond 3 months you cannot do it. So in this case, yes, it is fine. You're done. Okay, next one, the third one. Hey, I hope you're able to follow it quickly. I'm trying to do that so that you guys see different perceptions and different types of questions being asked on a topic which you guys would have already studied. Clear? Okay. Mr. Sohan, a wealthy individual, provided a loan of rupees 80,000 to Mr. Mukesh on 26th Feb 2023. The borrower, Mr. Mukesh, asked for further loan of 1,50,000. Mr. Sohan agreed but provided the loan in parts of different dates. That is 1,00,000 and 50,000. On 10th March, Mr. Mukesh, while paying off the part of 75,000, Mr. Sohan insisted that the lender should adjust 50,000 towards the loan taken on 3rd March and balance against the loan on 26th March. Mr. Sohan objected to his arrangement and asked the borrower adjust in order to date of, now you decide whether the contention of Mr. Mukesh correct or otherwise as per the provision of Indian Contract Act. Answer is yes, people. Appropriation of payment. The first option is always given to first option to the debtor. Second option, people, circumstances. Third option, people, creditor. Fourth option, people, first in, first out. Appropriation of payment, very important from exam point of view. What would be the answer in case borrower does not insist on order? Then it will be the order decided by the creditor. What would be the mode of adjustment or appropriation if neither creditor nor debtor insist? Then FIFO, first in, first out. That is in the order of first in, first out. Rama directs Shyam to sell laptops for him and agrees to give Shyam 11%. How many of you have watched the MTP series? In that this question was there. How many of you have watched? All of you have watched this question on MTP. So you tell me, logically, should I take up this question or should I say that, hey, go and watch it there? What do you want me to do? But yes, nonetheless, I'll do. Rama directs Shyam to sell laptops for him and agrees to give Shyam 11% commission on the sale price fixed by Rama for each laptop. As Government of India puts restriction on import of laptops, Rama thought that the prices of laptops might go up in near future and hence revokes Shyam's authority for any further sale. Shyam, before receiving the letter at his end, sold 5 laptops at the price fixed by Rama. Shyam asked for 11% commission on the sale of 5 laptops for rupee 1 lakh each. Explain under the provision of Indian Contract Act whether sale of laptops after revoking Shyam's authority is binding on Rama or not. Your Visha. I asked you whether you saw MTP or not. Did you see? Whether Shyam will be liable to recover his commission from Rama? If yes, what will be the amount of such commission? People, when will the agency be effectively revoked? Only when the agent is aware of it, he gets to know about it. So the answer is, people, yes, the agency has still not yet come to an end. You will be liable for whatever the agent has sold. What will be the commission? 1 laptop is 1 lakh. I've sold 5 laptops and the commission is 11%. I need to pay 55,000 as my commission. Rohan found a wallet in a restaurant. He inquired all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep the wallet safe. What is the case law? What is the case law? You guys have to remember the case law just like that. Which case law? Hallin versus Howler, the diamond case law. Whoever finds the lost goods will become the next to owner of the goods. So in this case, I will continue to be the owner. So the cashier cannot reject it. I have to get back the goods. So until the true owner is found, that I will only keep the goods. Paridhi, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer Mr. Mittal, owner of empty laptops, for purchase of laptop on credit amounting to 60,000 on 1st August 2022. She promised to pay back the outstanding amount with interest at 16% per annum. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Paridhi was asked to pay the outstanding amount with interest, she refused to pay, saying that she is a minor. She will be a major on 1st January and only after that agreement can be ratified. Explain by which of the following ways Mr. Vittal will succeed in recovering the amount. By filing a case against Paridhi, a minor, for recovery of outstanding. Will he? Answer is no. Mohari Bibi versus Dharmodas Ghosh. Any minor agreement is void ab initio. By filing a case against Mr. Ram, father of Paridhi, for recovery of outstanding amount. Minor cannot bind guardians, so the father or the parents will not be liable. By filing a case against Paridhi, a minor, for recovery of outstanding amount after she attains majority, minor agreements cannot be ratified. So in none of the case the person will succeed. State with reasons whether the following agreements are valid or void. Where two courts have jurisdiction to try a suit, an agreement between the parties that the suit should be filed in one of those courts and not in the other. It is a valid contract. It is not agreement in restraint of legal proceedings. I am allowing you to file, but in the two courts you have to file a case on one. You have to go to one court, not the other court. Such agreement is valid or invalid? It is still valid only. It is valid. Next one. X offers to sell his Maruti car to Y. Y believes that X has only WagonR. People, bilateral mistake, void agreement. X a physician, a mistake of fact, subject matter. X a physician and surgeon employs Y as an assistant on a salary of 75,000 per month for a term of 2 years, and Y agrees not to practice as a surgeon and physician during these 2 years. As an employee, people, agreement in restraint of trade, business, profession, as long as your employee is valid, hence it's a valid agreement. R owns an electronics store. P visited the store to buy a water purifier priced at 54,000. He specifically requested R for a purifier with a copper filter. This I have done it in MTP. I am telling you guys to go and watch it this time. Watch it. Yeah. What are the conditions? Okay, this is done direct. Let us not do. Shubhangi went to a jewelry shop and asked the sales girl to show her a diamond necklace with sapphire stones. The sapphire song. The jeweler told her that we have a lot of designs of diamond necklace but with the blue stones. If she chooses for herself any special design of diamond necklace with blue stone, they will replace the blue stone with sapphire stones. But for sapphire stone, they will charge some extra cost. Shubhangi selected a beautiful designer necklace and paid for it. She also paid the extra cost for sapphire stones. The jeweler requested her to come back a week later for delivery of that necklace. When she came back after a week to take delivery of necklace, she noticed that due to sapphire stones, the design of necklace had been completely disturbed. Now she wants to terminate the contract. Thus asked the manager to give her money back. So state with reasons whether Shubhangi can recover. Answer is yes, she can recover. Because the condition is clear that this is what is my condition. The condition is not met. Quality of fitness does not suit my purpose. What would be your answer if jeweler says that he can change the design but he will charge extra cost? He cannot charge the money, people. It is your duty to make good the default. So you cannot charge for it. Yes. J, a wholesaler of premium basmati rice, delivered on approval 100 bags of rice of 10 kg each to a local retailer on sale or returnable basis within a month of delivery. The next day, the retailer sold 5 bags to a rice of regular customer. Again, we have done this in MTP, requesting you to watch it once. Mr. Kanchan, MTP, it is done. Watch it once. Clear? Because we have done it again, same thing. Why repeat? New questions will take it up. Ravi sold 500 bags of wheat. People, but what do you guys think? Is this helping you? Is it not helping you? Question number 1. Question number 2. What more you think you need to give a confident attempt? And tomorrow again, I'm telling you, we are doing the writing practice. Apart from that, what more you think you need to write a confident attempt? You put it in the comment section below. And by the way, I hope you know that I gave you, a lot of people were asking me, sir, give us your chart book. And I gave the chart book also to you. If you guys have missed it, just go and see in this mission 80, the second day we have uploaded the chart book. In our first day in the marathon itself, the chart book is made available. So go and get your chart books if you guys want it. Yes, and it's free. But what else you want, you let me know. Ravi sold 500 bags of wheat to Tushar. Each bag contains 50 kgs of wheat. Ravi sent 450 bags by road and Tushar himself took remaining 50 bags. Before Tushar receives delivery of 450 bags sent by road transport, he becomes bankrupt. Ravi, being still unpaid, stops the bag in transit. The official receiver on Tushar's insolvency claims that the bags cannot be stopped. Decide the case. People, whatever is delivered, the 50 kgs, I cannot do anything on it. Whatever is the 450 kg which is on the way, it is still in a transit. Because it is still on the way, it is not yet reached. On that, can I exercise my right to stoppage in transit? Answer is yes. So the total contracted quantity was 500 kgs or 500 bags. In that 50 is delivered. Once delivered, on that I do not have stoppage in transit. For whatever is not delivered, I can exercise the right to stoppage in transit. See, that is how you need to write your provision. I can exercise right to stoppage in transit. Clear? Okay, direct. PQ and R formed a partnership agreement to operate motor buses along specific routes for a duration of 12 years. MTP. What is this? Perpetual losses. What can you do? You can go to the court asking for dissolution if there is a perpetual losses. That's the answer. Ram and Shyam are partners in a partnership firm styled as RS & Co. Gopal, a renowned businessman, is their common friend. MTP. What is this? Partner by holding out. At least for this, you guys will go and watch. Go and watch. Partner by holding out. Next one, company. BC Private Limited and its subsidiary KL Private Limited are holding 90 and 70,000 shares respectively in PQ Limited. See how I will write a subsidiary company. BC and KL are holding PQ in PQ. They are holding 90,000, 70,000 shares. The paid up share capital of PQ is people 30 lakhs. That is 3 lakh shares. The total they have is 3 lakh. How much are they together holding? 1.6 lakh together they are holding. Okay. Analyze with reference to the provision of Companies Act whether PQ Private Limited is a subsidiary of BC Private Limited. Okay, BC Private Limited and its subsidiary KL. So KL is its subsidiary. Then yes, people, of course, PQ is a deemed subsidiary of BC. Of course. What would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC Private Limited? So what if 90 is not held? Directly KL is holding 1.6 it seems. Even then, people, it is a subsidiary, deemed subsidiary company. It is this order. It is still a deemed subsidiary. Narendra Motors Limited is a government company. Shah Auto Private Limited have share capital of 10 crore in the form of 10 lakh shares of 100 each. Narendra Motor Limited is holding 5 lakh 5,000 shares in Shah Auto Private Limited. 5 lakh 5,000, that is more than 51%. Is it a government company? Of course, it is a government company. XYZ company incorporated under the Companies Act 2013. The paid up share capital of XYZ. Government of India is 20. I will not count 8%. I will count Government of Tamil Nadu. 20 plus 10, 30. I'll count Rajasthan, 40. I'll not count this. So I'm only holding 40%. So is it a government company? Answer is no. Mr. Y issued a check for 10,000 to Z which was dishonored. MTP. What is the consequence of dishonor of a checkda? Imprisonment of 2 years or fine up to 2 times of the amount of the check or both. So amount of check is 10,000. The penalty can go up to 20,000. Reliable Limited, an Indian company, is a global leader in petrochemical products. For payment of the sale price of machinery imported from again MTP. See, I'm telling you, see the commonalities. Yeah. So this is nothing but a question on inland instrument. Now the question for you, when will a instrument be considered as inland instrument? When the instrument is drafted, drawn in India, payable in India, or drawee resides in India. So drawn in India and payable in India or drawee resides in India. So this condition mandatory. In these two conditions, any one, then it is a inland instrument. Done. Next one, Sri Shivai Temple Trust decided to get renovation of the temple under trust. For this purpose, the president of trust discussed the budget. Again, people, MTP. What is this, people? This is nothing but charity, quid pro quo, exception to quid pro quo, people, charity. So when one person promises to pay another person some money as a charity, is it a valid contract? Yes, provided if the person has undertaken any liability. Case law you can quote here, Kedarnath versus Gori Mohammed. Yeah. Sahil deals in pre-owned cars. Raju sold his accidental car to Sahil by fraud. My God. Sahil could not find that the car was accidental. So Sahil sold it to Raju. No. Raju sold it to Sahil. And Sahil further sold it to Akshay. This was fraud. Akshay informed Sahil his intention with condition that car should be free from any accident. Sahil sold that car to Akshay on erroneously believing that the car did not face any accident. Afterwards, Akshay found that the car was actually an accidental case. He sued Sahil to avoid the contract and also for damages for expenses suffered on car. Taking into account the provision of Indian Contract Act, state whether Akshay was eligible to avoid this contract. The answer is yes, people. This is misrepresentation. Because Sahil was also not aware that the car was, a accident car. Even Sahil was also not aware of it. Hence, the Sahil sold to, Akshay, thinking that the car is fine because he thought it is fine. So it's a misrepresentation. Can I avoid the contract? Yes, the contract is voidable, but you are not eligible for any compensation. Compensation will come into picture only if fraud is involved. Yes, I can avoid the contract. Rahul is manufacturer of jute bags. He contracted with Sonia to supply raw jute for the purpose of making bags. Rahul informed Sonia that production process of jute bags would start from 27th June. But Sonia must supply the raw jute on 25th June so that the quality verifications can be done in the next 2 days. Sonia supplied the jute on 27th June only. Breach of contract. And informed Rahul that she couldn't supply on 25th June due to some unavoidable reason, and she also assured that the quality measures were not anyway compromised in supplies. But Rahul wanted to avoid the contract as he was not given opportunity to examine the goods. In light of the Indian Contract Act, whether Rahul can avoid? Answer is yes. Breach of contract, failure to perform within the reasonable time. When time is essential, I can avoid the contract and hence the contract is void. It can be considered as void. You can cancel, you can rescind the contract. Mr. Janta Machine Tools and Company contracted with Measures Ruchi Traders to make and deliver certain machinery by 31st July for 15 lakh. There was a labor strike in the factory of Measures Janta Machine Tools and Co. and it could not manufacture and deliver the machinery to Measures Ruchi Traders. It was a labor strike. Okay. Afterwards, Ruchi Traders had to purchase the machinery from another manufacturer for 18 lakh. Measures Ruchi Traders was also prevented from performing a contract which was made with Measures Shiksha Technologies at the time of the contract with Measures Janta Machinery Tools, and company were compelled to pay compensation of 2 lakh to Measures Shiksha Technologies. Measures Janta Machineries, Machine Tools and Co. was very well informed by Measures Ruchi Traders about its contract. I can recover ordinary damages also. I can recover special damages also because the special circumstance was communicated. I've told that there is an ongoing contract. So even after telling them, if you do not, I can recover special damages. Ankit has taken a loan of 1 lakh from Kishore on the guarantee of Sudeep at the interest of the rate of 12%. After some time, due to financial crisis and at his request, Kishore reduced the rate of interest to 8% and also extended the time of repayment of loan without the consent of Sudeep. Ankit becomes insolvent. Whether Kishore sue Sudeep for recovery of the amount under the provision of no people, surety will be discharged if there is any variation in the contract. Ram Billas Yadav is a farmer. Anna Chips company approached him and entered in a contract to supply 100 quintals of potatoes, which to be grown in the fields belonging to Ram Billas Yadav at 1000 per quintal. Anna Chips company made the payment of price, but delivery to be made after 6 months. Okay, they have entered into a contract today, but delivery in the future. Before the time of delivery, the whole crop of the potatoes were destroyed due to flood. Anna Chips company demanded the payment of price which it already made by it. Ram Billas Yadav denied retaining the price by saying that the contract of sale was already entered and hence crop belonging to Anna Chips company, hence loss of crop must be borne by it. Referring people, remember, it's a agreement to sell. It's a future goods. The ownership will not transfer until the goods are future goods. So until it is produced and until it is ascertained, the ownership will not pass. So here the ownership will always be on the farmer only. So the risk will be on the farmer. Kapil entered into a contract with Rahul to purchase 1000 liters of mustard oil at the price which should be fixed by Akhilesh. Rahul already delivered 600 liters out of 1000 to Kapil, but remaining 400 was ready to deliver. Akhilesh denied fixing the price of mustard oil. Rahul asked Kapil to return the oil already delivered and avoid the delivery of 400 liters. Kapil sued Rahul for non-delivery of remaining 400 liters. Advice in the light of Sale of Goods Act. People, whenever we have appointed a valuer to come up with a valuation, if the person is not able to arrive at a number, price, then we can avoid such contracts. We can set aside that contract. But however, if at all the goods are already delivered, if you have already given the goods, in such case, what will happen, people? If the goods are already delivered, correct? If the goods are already delivered, what will happen in such case? In such case, people, reasonable price should be paid for 600. This cannot be cancelled. 400 can be avoided. Saurabh purchased electric scooter of Vivek for 5,000 only on the gunpoint. Vivek decided to file the complaint and to avoid the contract on the basis of coercion applied against him by Saurabh. But before he could do that, Saurabh sold the scooter to Vinay, who had no idea about the situation on which the scooter was purchased by Saurabh. Vivek sued Saurabh and Vinay for recovery of scooter, referring to the provision of Sale of Goods Act, whether Vivek was correct in his decision. People, sale of goods by a non-owner, nemo dat quod non habet, exceptions to that. A person in possession under voidable contract, the ownership can be properly passed. If the contract is not yet cancelled or rescinded, the ownership can be passed, and hence, people, it is a valid contract. Amit and Ajay started the business of wholesale trading the sugar For this purpose, they contributed 3 lakh and 1 lakh respectively. Partnership deed was perfectly prepared, but clause regarding the share of profit was not mentioned in the deed. Due to heavy rain, the stock of sugar was spoiled and firm incurred the loss of 60,000. Amit asked Ajay to contribute equally, but Ajay agreed to contribute only 25% of the loss in the ratio of capital. People, the profits and losses will always be distributed as per the ratio agreed by the partners in the agreement. If the agreement is silent, people, it will always be distributed equally, not in the profit, not in the capital ratio. So it is equally clear. So it will be equal. Yes. What is the difference between, okay, state giving reasons whether the following are partnerships or not. XYZ agree to divide the profits equally, but the loss, if any, is to be borne by X alone. Is it valid? Yes. Profits has to be mandatorily shared. Loss can be taken by one partner. It is allowed. It is okay. It is still a valid partnership. X, a publisher, agrees to publish a book at his own expense written by Y and to pay Y half of the net profit. Does this create a relationship of partnership between X and Y? X, a publisher, agrees to publish a book at his own expense written by Y. Okay, 1 second. Flickering is happening. Huh? Huh. Agrees to publish his book at his own expense written and by Y and to pay Y half of the net profit. Now, does this create a relationship of partnership between X and Y? So people, let us take a business is done by him, book at his own expense written by Y and to pay Y half of the net profit. People, you are just sharing like an interest, people. There is no business. There is no mutual agency. There is nothing. So I cannot call it as a partnership. Current is going. A and B purchase a tea shop and incur additional expense for purchasing utensils, each contributing half of the total expense. The shop is leased out on daily rent, which is divided between both. Does this arrangement constitute a partnership? Of course, no. It's a lease. Are they doing business? Answer is no. They're just giving it out and someone else is doing the business. So is it a partnership? No business is happening. Ratan Mul Milk India Limited is a public company and formed on on this day Mr. Sharman was appointed as legal advisor of the company. It was mentioned in the articles of the company that Mr. Sharman will not be removed from the post of legal advisor till 31st March 2027. On 1st July 2024, a special resolution was passed for the alteration in the articles and Mr. Sharman was removed from the company. Mr. Sharman filed a suit against Ratan Mul for removal as legal advisor. Whether can company remove Mr. Sharman? People, remember people, articles of association is always an internal document. Legal advisor is an outsider. It will never bind the outsider to the company. It is always for the shareholders. This particular articles are there. Anything written in articles, people, it does not create any contract between company and an outsider. So in our case, people, it will not bind the legal advisor to the company. So can we remove him? Yes, we are free to remove because it is written in articles of association. It does not create a contract with him. So we can remove. XYZ was incorporated to hold MTP, dormant company. It cannot be a dormant company because they have invested 1 crore. Go through the question. There is a significant accounting transaction. So it cannot be a dormant company. Priyansh purchased some goods from Sumit. He issued a check to Sumit for sale price. Sumit presented the check in his bank and his bank informed him on 19th June. Just now we saw dishonor of a check. A promissory note payable at certain price. Done. Last one, people. Taka will do. Come on. Albert obtained 2 loans of 3 lakh and 4 lakh respectively. People, again, we just did appropriation of payment. Okay, CS Sarthak Jain has decided to get interior work for his new office. For this purpose, he entered into a contract with Measures Sharif Fine Interiors. It was agreed that Measures Sharif Fine Interiors will complete the interior work up to 31st Jan 2025. On 31st Jan 2025, CS Sarthak Jain observed that only 20 to 30% work is completed. He decided to cancel the contract with Measures Sharif Fine Interiors. Sharif Fine Interiors filed a suit against the CS Sarthak Jain for recovery of the cost which he incurred on the interior work. CS Sarthak Jain argued that Sharif Fine Interiors did not complete the work within the time, and further the work done was of no use to him as he has to appoint a new interior designer. Explain whether CS Sarthak Jain is liable to pay the cost of work done. People, they are trying to confuse you with the quantum merit. But remember, this word plays a very major role. Which word? This one. If the 20-30 percentage, if it is of any use, then yes, I cannot say that I'll deduct you complete money and I'll not even give you 1 rupee. I cannot say that. But in our case, people, what has happened? In our case, whatever work you have done is absolutely unfit. I have to get everything redone. Literally everything is to be done from the scratch. In such case, whatever you have done, what is the use? So, can I cancel the contract? Yes. Should I pay some money? Absolutely no. Is clear? Done. Rohan of 17 years has purchased a mobile of 25,000 for his online classes from Mobile Sales Center on credit. Online classes. Education. On the due date, he did not make the payment of mobile. Mobile Sales Center sued Rohan and his parents. Minor cannot bind guardians. Rohan has 15,000 as his cash balance, but his father has enough money to pay the price. Examine the given situation. Minor will be liable for necessities, education. So whatever is my asset to the extent of 15,000, I will be liable. Akhil ordered 100 kgs of wheat to Measure Sahil Kirana store and it promised to supply the wheat by the evening. In the evening, the hawker of Measure Sahil Kirana store comes with, meaning dealer, with 100 kgs of wheat, but mistakenly he delivered it at the house of the neighbor of Akhil. Referring to the provisions of Indian Contract Act, advise who will be liable to pay the price of the wheat. People, quasi-contract people, any person who has taken the benefit under mistake, you will have to repay it. Quasi-contract. So the neighbor has to pay the money. You don't have a choice. Rahul hired a car for 15 days from Measures Kushwa Travelers. After 5 days, Measures Kushwa Travelers demanded back his car. See, contract was entered for 15 days. They have asked back after 5 days. And people, it is hired. That is for money. So you don't even have to see the next part of the question. Whenever it is bailment, hire is a bailment only, no? Two types of bailment can happen. One is gratuitous, non-gratuitous. Non-gratuitous means, people, whenever bailment for money, for hire, such bailments, people, you cannot cancel it before the scheduled time. So in this case, you cannot cancel it as long as they have not done a misappropriation of goods. So in this case, no, you cannot cancel because it is a bailment for hire. Ajay appoints Vijay to sell his electronic goods lying in his godown. He also agrees to give 10% commission on sale price to Vijay. Afterwards, Ajay revokes Vijay's authority by sending the letter to Vijay. Revocation of agency. When will it be effective? Whenever the agent gets to know. That laptop, same thing. Mr. G sold some goods to Mr. H for a certain price by issue of an invoice, but payment in respect to the same was not received on that day. The goods were packed and lying in the godown of Mr. G. The goods were inspected by H's agent and were found to be in order. Later on the day, dues, the goods were settled in cash. Just after receiving cash, Mr. G asked Mr. H that goods should be taken away from his godown to enable him to store other goods purchased by him. After one day, since Mr. H did not take delivery of goods, G kept the goods out of the godown in open space. Due to rain, the goods were damaged. Who will bear the loss? People, when does the ownership transfer? Risk prima facie transfers with the ownership. So people, delivery and price is irrespective, people. Once the goods are ascertained, appropriated, the ownership transfers. But people, remember the seller's duty as a bailee to keep the goods safe. You are always liable. But provided he took a reasonable care of the goods, but he had to keep it outside because he had to keep some other goods inside. So because of that, I kept outside. So will I be liable for that? No. As a bailee, I have taken proper care of the goods. So who will be liable? People, the buyer will be liable. The seller will not be liable. Measure CMA 125 kg MTP. We saw it today also. Raghav arranges an auction to sell an antique wall clock. Deepa, being one of the bidders, gives the highest bid for announcing the completion of sale. The auctioneer falls the hammer on table, but suddenly hammer breaks and damages the clock only. People, in auction, people, when does the ownership pass? When the hammer hits the table 3 times or whatever is the customary. Here it is not yet done. So people, the sale is not yet done. So the seller will only be liable, not the buyer, because the sale has not yet happened. X contracted to sell his car to Y. They did not discuss the price. What is it, people? Reasonable price is to be paid. A and B are partners in measures A, B and company. Firm is doing business of trading of plastic bottles. A is authorized to sell the stock of plastic bottles. It was decided between them that A should sell the plastic bottles at a minimum price which they have decided, and if A sells at a price less than the minimum price, he should first take the permission of B. Due to sudden change in government policy, the price of plastic bottles was continuously declining. To save the loss of the firm, A sold the stock at a lower price. Meanwhile, A tried to contact B but could not do so as B was on a foreign trip. Afterwards, B came and filed a suit to recover the different sale price and minimum price of the firm. Whether B can do so under provision. Indian Partnership Act, people, answer is no. Partner can sell or can go even beyond his authority during the necessity. So here the commercial necessity, I tried calling you, you were not reachable. In such case, what do? B cannot recover because partnership by necessity, I can do anything, you are liable. Done. Ram and Rahim, Ishwar Chand, we just did today only. Not even RTP, today only we did it. PQ and R formed a partnership agreement, 12 years, people. Perpetual losses, MTP, we have done this. A and B operate a textile merchant business in partnership. Mr. A finances the business and is a sleeping partner. MTP, we have done this. Tycoon Private Limited, again we have done this. MTP, watch it. In the Flower Fans Private Limited, there are only 5 members. All of them went on a pleasure trip. Again, we have done it. What is this, people? 5 shareholders go on a trip, da. All of them die. Will company come to an end, da? No, perpetual succession. The legal heirs will continue the business. An employee, Mr. Karan, signed a contract with his employer company that he will not solicit the customers after leaving the employment from the company. Today only we did Clifford Motor Company versus Horn. Pacific Motors Limited is a government company. Rama Auto Private Limited is a private company having share capital 10 crore in the, just now, today only we did it. A subsidiary of a government company is a deemed government company. See, that's why I say questions will repeat. That's why I say now, see, you see 5 MTPs, 5 RTPs. It's like seeing 10 question papers, da. See, the questions are repeating, no. Getting my point? Yeah. Aman drew the bill on Baban, MTP. We have done this. Reliable Limited. Today only we did. Is it an inland instrument or a foreign instrument? It's an inland instrument. Done. Dana. Macha Danda. 5 RTPs. People. So let me know if you guys want to see anything else. You want any other support. But make sure you guys make it count in law. Tomorrow I will be presenting how to present the answer. I will write and show. Yeah, sir, will you write only one answer? No, I'll write 2, 3. How many you want me to write? We'll write at least 3 answers. We'll at least write by practicing 3 answers. So even I'll try to become a student. We'll see how I will write. And you also see. And see, let us learn something out of it. Apart from this, if you guys want something else, do let me know. Yes. So thank you so much for today. Let us meet tomorrow session. See you all people. Bye-bye. Hello guys. I hope you guys are doing good, and you guys have completed our last 3 days of sessions as per our schedule. Marathons, I hope you guys have watched, and I hope you have seen the most important topics, and you have also covered the case laws. They please go and see the That's the least we can do. Yes or no? At least make the maximum utilization of all those resources. Yeah. So today's agenda, people, let us solve at least 5 MTPs. See, good enough. At least in one paper, 20 questions, 22 questions will be there. So sit back and relax. Wherever you guys know the answer, pause it and you only try to tell. And then see the solution, what I'll be telling. See if there is a match. By that you will be, end of the day, in this whatever the video duration, you'll be able to cover 100 questions. No, good, right? Okay, let's start. So we are doing 5 MTPs for today, and that will be the agenda. Tomorrow it will be 5 RTPs. Yep. Okay, so let's start. PQR jointly promised to pay S a sum of 60,000. Examine considering the provisions of Indian Contract Act 1872. Can S compel any of the 3 parties P, Q and R to pay him 60,000? Is it possible? Answer is yes, it is possible. Remember, joint promisors is one of the important topics. In our most important topics, I have put this also. So whenever there are 3 joint promisors, can the promisee, that is, imagine if there is a creditor, can he recover money from any one of the person? The answer is yes. Now imagine, can I compel, can S compel any of the 3 parties? Imagine, can I compel P alone? Yes, you can compel, but P can later on recover it from Q and R. Possible. R is compelled to pay the whole of the amount. R is compelled to pay it seems. Okay. To S, can he recover from P and Q? Yes, possible. Agreed? Oh, they have given sub scenarios. When both P and Q are solvents, when they have money, of course you can recover. P is not in a position to pay anything, meaning let us imagine P has become insolvent. When you have become insolvent, people, then I cannot recover. In such case, what will happen? Q and R have to bear the loss, so you need to pay 30,000 each. Try to show this number and put it in your exam. Instead of just saying that whether you can recover, you cannot recover, tell them how much you can recover, how much you cannot recover. Be very specific. Getting the point? Now here I am just discussing the solutions. I am not discussing how to write and all. Day after tomorrow, that's the last day of our Mission 80 series. The last day, people will be seeing on how to present it. Now I'll be taking up these questions and I'll also try to write along with you. Try to learn how to write that time. Yep. Now let us focus on solving more and more questions inside the class. Okay, because remember, the key for your law is, people, the more questions you see. Second one is the art of writing. You need to get these 2. Okay, next one, Oakwood Private Limited is a holding company of Silver Oak Private Limited. Okay, Oat is a holding company of Silver Oak. As per the last profit and loss account for the year ending of Silver Oak Private Limited, its turnover is 1.8 crore. Its turnover is 1.8 crore and paid up capital is 80 lakh. The board wants to avail the status of small company. Possible. A CS, the company advised the Silver Oak cannot be categorized. Please give your possible people. What is small company, people? As per section 2 clause 85. A company other than public company whose paid up capital does not exceed 4 crore, turnover does not exceed 40 crore. But it does not include holding, subsidiary, statutory and Section 8 company. Silver Oak is a subsidiary company and hence Silver Oak cannot be categorized as what? It cannot be categorized a small company. So yes, company secretary's contention is valid. In the Blossom Private Limited, there are only 5 members, all of them going in a boat on a pleasure trip into a open sea. The boat capsizes and all of them died being drowned. My God. Explain with reference to the provision of Companies Act. People, what are they trying to tell you? They are talking about people perpetual succession. So once a company is a separate legal entity, perpetual succession, members may come, members may go, but the company will go on forever. So in this case, the legal heirs will get the right to carry out the company. Is it no longer in existence? No, it will continue to be in existence because it's a perpetual succession. Is it correct to say that a company being an artificial person cannot own property and cannot sue or be sued? No, this is incorrect. A company is an artificial person and recognized as a body corporate in the eyes of the law, and hence it is eligible to hold property in its name, can sue, be sued. Explain the rules laid down under Indian Partnership Act for the mode of settlement of partnership accounts after dissolution of what is the order in which assets of the firms are applied. How it is, first people, losses if any, mode of settlement of partnership accounts after dissolution of a firm. So what do we do? First we will repay third parties debts. Next, loans and advances, anything over and above capital, and then capital, and anything surplus will be distributed. Discuss the provision of Indian Partnership Act regarding the payment of firm's debts and separate debts. The firm's properties will be used to first repay the firm's debt and then separate debt. Whereas on the other end, the separate debt of the partners will be used to first repay the separate debt of the partners, and if there is still excess, then it will be used to repay the firm's debt. Correct? Done. The Institute of Science and Technology, Dehradun, placed an order for various chemicals worth 1,50,000 from a supplier in Delhi. The buyer made full advance payment and the seller dispatched the consignment via courier of his own choice without reserving any right of disposal over the goods. The consignment was lost in transit, and now the buyer seeks a refund for the purchase of the price. With reference to the provision of Sale of Goods Act, when does the ownership pass? People remember, when does the ownership pass? Whenever the goods are given to a courier, whenever the goods are given to a carrier, and if the goods are ascertained and unconditionally appropriated, and there is no right of disposal reserved. So if at all that carrier, the courier, if he is appointed by the seller or not, if the goods are given to him, then the goods are considered as if it's unconditionally appropriated. So the ownership passes people the moment it is given to that person. So because the goods are given, so A is selling some goods to B by a courier. It is shipped by a courier. People remember, payment and delivery is irrespective. If the goods are appropriated and if it is clearly given without reserving a right of disposal, people, that's all it's done. The goods are appropriated. The ownership is passed. So can you recover the loss? Answer is no. Siddharth visited an authorized car showroom and purchased the car of his own choice without conducting a detailed inspection. After making the payment and taking delivery of the car, he discovered a defect in the engine that could not have been detected even with a reasonable inspection. With reference to the provisions of Sale of Goods Act, advise whether Siddharth can invoke the implied condition of merchantability and repudiate the contract due to the defect in a car. Yes, people, possible, because these are called as what people, latent mistakes, we call it. Meaning even if you check, if you cannot identify it, we call them as people hidden or latent mistakes. So such things, people, yes, you can invoke the implied condition as to merchantability. What do you mean by merchantability? The product that you are buying, people, should always be free from defects. Yes, can I? Yes, I can. Agreed. Explain the classification of capital. What is the authorized capital? Issued capital, subscribed capital, called up capital, paid up capital, that one. Direct ones, let us not go through. Explain advantages of LLP form of business. Whatever you write for company, write the same thing, it will still be valid. P, Q and R are the partners in a construction firm. P, Q are associates. P buys the cement on behalf of the firm from D. The cement is used in the ordinary course of the firm's business. P uses the cement for his personal purpose. The supplier D, who is unaware of the private use of the cement by P, claims the price from the firm. The firm refuses to pay for the price on the ground that the cement was never received by it. Referring to the provisions, answer whether the firm's contention is tenable. What would be your answer if a part of the cement so purchased by P was delivered to the firm by him and the rest of the cement was used by him for his private purpose, about which neither the firm nor the supplier were aware? So what is happening, people? One partner takes cement and cement is used by the partnership firm in the ordinary course of business. So remember, a partnership firm will always be liable if the goods are purchased or if any contract is entered by any partner in the ordinary course of business, meaning cement is their everyday activity. Second one, people, the partner should have acted within his authority, within the scope. In such case, any contract entered by P, the firm will be liable provided if that particular contract was entered in the name of the firm. So P has clearly said, I am a partner in PQR firm, I am borrowing this cement for the firm. So in this case, people, whether P, Q, R, will they be liable? Yes, people, the firm is liable. Mutual agency. Agreed? Yes. Sir, what if half was given to the firm and half he used it? Even otherwise, you are liable for the full thing only. If that particular cement was purchased in the name of the firm in the ordinary course of business, the firm will be liable. Any misappropriation will not stop the liability of the firm. Firm will be liable. Later on, can I file a case on P? Yes, sir. Amongst you guys, you can file a case. But you cannot file a case or you cannot exclude your liability from the third party. Unity Foundation is a newly incorporated company focused on promoting education and healthcare services in rural areas. The company is registered as Section 8 company. It's a Section 8 company. Okay. With a clear plan to reinvest all profits into activities. Very good. And the license has been accorded by the central government. Very good. For the financial year, the company earned a substantial profit and transferred some amount to measures ABC Associates, a partnership firm, and one of the member in that particular Section 8 company. Okay, they have transferred some profits to a partnership firm which is a member in this particular company, it seems. Remember, only exception. A Section 8 company can become a member in, a partnership firm can become a member in Section 8 company, or else generally partnership firm cannot become a shareholder. Only exception is Section 8 company. And transferred some amount to measure, okay. Subsequently, on the complaint of one of the members, the central government, after giving an opportunity of being heard, directed the company to be wound up. That a partnership firm cannot be a member of Section 8 company and it cannot transfer any part of the profit to the firm. Explain the right of the provisions of Companies Act. People, what has happened here, people? There is a Section 8 company. In this Section 8 company, there is a shareholder and that shareholder is a partnership firm. First problem they have is, can a partnership firm be a shareholder in a company? Answer is yes, we don't have a problem. On this, you cannot wind up that partnership. You cannot wind up a Section 8 company. This is not any non-compliance. It is in proper compliance only. Second one, people, can a Section 8 company give any part of its profits to any person? Forget about partnership. Can you give it to any person? No, people. Distribution of dividend is always prohibited in a Section 8 company. On this ground, people, the Section 8 company has done a violation. So central government may pass an order if it deems fit. Yes, the central government's order will be valid. Simple. Okay. Pacific Private Limited has 9 directors on its board. The company's articles of associations currently state that the quorum for board meeting is 1/3 of the total strength or 2 directors, whichever is higher. The company now intends to amend this article to specify that The quorum for board meeting shall be 1/3 of the total strength or 4 directors, whichever is higher. Currently it is 1/3 or 2, whichever is higher. They want to make it 1/3 or 4, whichever is higher. Possible? Yes, people. Remember, this is only called as nothing but, yes, what? Section 5, people. Entrenchment of articles of association. If at all, people, okay, it's a Pacific Private Limited. How can a private company entrench its articles of association? By passing a resolution which is accepted by all the members. All the shareholders have to agree. Would your answer be different if the company is public company? Yes, my answer will be different. If at all it is a public company, for the entrenchment of articles, special resolution has to be passed. Once it is passed, kindly intimate ROC, and then yes, this particular changes will take place. Is clear, all of you? And the provision they're asking you people is on entrenchment of articles. If you guys remember, see, in the most important topics, all this I have told you to study. Entrenchment and all. Don't leave it. What is an anticipatory breach? Before the due date, if the contract is called off, anticipatory breach. Okay. Examine the validity of the following agreements under the Indian Contract Act. Ms. Deepika pays a sum of 20,000 to a marriage bureau to provide information. Is it opposed to public policy? No, people. It is absolutely valid. Remember, marriage brokerage agreements are different from marriage bureaus. They do not do a brokerage. They just sell you the data. So this agreement, this contract is valid. Bharat agrees with Rahul to sell his white horse. Unknown to both the parties, the horse was dead at the time of agreement. Mistake of fact. Both of them did not know. So bilateral mistake of fact. Bilateral mistake, the contract will always become, it's a void agreement. Agreed? Next one. Ayush sells the goodwill of his shop to Omkar for 5 lakh rupees and promises not to carry on such similar business within the local limits so long as Omkar carries on like business. Meaning, sir, A sold his business to B and clearly said that B is telling people, I will buy provided you cannot start a similar business in the same local area. Is this restriction valid? Answer is yes, people. Restriction in, restriction in trade, it will be valid provided people, the restriction is always reasonable. If it is unreasonable, people, then no, restrictions cannot be, it will not be valid. So in this case, what are they telling you? They're telling you cannot carry on a competing business in the local area. What if I can go a little far and can I do? Yes, I can do. They are not restricting me forever or from everywhere. It is only from a particular place. It is valid. A property worth 20 lakh was agreed to be sold for just 2,50,000 by a person of unsound mind. People will just, in rush, they will write off the answer. Sir, the consideration may be inadequate. They will just write that and they'll come off. People remember, unsound mind, the contract of course is invalid. What is negotiable instrument and its characteristics? I think manageable. RBIC, remember and go. MCA, remember and go. Okay. PQR Limited, a supplier of electronic components, entered into a contract on August 1st, 2024 with PQR Enterprises for a sale of 1,000 units of microchips. The contract specifically identified the microchips by serial numbers. So see, what do you mean by that? Amongst the bulk, what they want is already ascertained. So the goods are identified. That means ownership should have been passed. And confirm that they were in the deliverable state. So goods are also in deliverable state and identified. Specific goods. So the contract is made. Ownership is passed whenever the contract is made. Stored in PQR Limited's warehouse. The contract stipulated that the goods would be delivered on September 1st, 2024. Contract is entered on 1st August 2024. So people, I'll tell you, will not even read the question. If at all the goods are in deliverable state and if at all the goods are ascertained and if the goods are appropriated, meaning selected, everything is done. In such case, people, the ownership passes immediately. The payment of price and the delivery of goods are irrelevant. So people, the ownership passed on August 1st only. Anything happens after August 1st, people, the liability will be on the buyer, not on the seller. That's what they are. See, on August 10th, flood occurred, damaged the warehouse, destroyed the entire stock. In such case, who will be liable? Buyer only will be liable. Ownership is passed. Done. A purchases a motorcycle from B and uses it for some time. It turns out that the motorcycle sold by A to B to A was stolen one and had to be returned to a rightful owner. A brings action against B for the return of the price. Will this person succeed? Implied condition as to the title, people. If at all A sold the goods to B, we assume that A is the owner. What if it was a stolen goods? Then people, B will have to return the stolen goods to the actual owner. Whoever is the actual owner, you have to transfer it to them. And later B can recover the money from A. This is possible. Is the answer possible? Yes, possible. You can recover the price. Done. What is partnership deed? Enumerate obligation. Yeah, okay. Kanika purchased various cosmetic products worth 15,000 during the last week from Karthik, a shopkeeper, on credit of 1 month. After a fortnight, she makes out a blank promissory note, signed it, and delivered it to Karthik, who further endorsed it to Manish. Kanika gave a promissory note to Karthik. So she has to make the payment. Okay, what is Karthik doing? Karthik further endorsed it to Manish for the payment of his dues. Manish, who is a holder in due course, Manish is HDC Sims, holder in due course, filled up the due amount of 17,000. The actual value of Kanika given is 15,000. What Manish has filled in it's a blank instrument, no? They have said no. Blank promissory note. Manish filled 17,000. And her maturity presented to Kanika for payment, but she refused to pay because the amount filled up is more than the agreed amount, 15,000. It is to be noted that the amount of 17,000 is covered by the stamp affixed on it. Referring to the provisions of Negotiable Instrument Act, whether Kanika is liable to honor the promissory note to Manish for 70,000. Yes, people, always remember, if you are a holder in due course, you are eligible to recover whatever is the money up to which the stamp duty is covered. Correct? Yes, sir. So, sir, if Karthik had to pay Manish 17,000, if Karthik owes Manish 17,000 and the stamp duty also covers it, people, then yes, I will be liable. I can recover the entire 17,000. Kanika cannot say that I am responsible only for 15,000. Yes, sir, I can recover up to the stamp duty covered. Okay. Nisha, a small business owner, receives a bill of exchange from her customer Neeraj, which is due for payment on October 15th. On October 12th, Nisha presents the bill of exchange for presentment at Neeraj's office during business hours. But Neeraj is not present. Nisha leaves the bill with Neeraj's assistance, requiring to be presented to Neeraj for payment when he turns. However, Neeraj's assistants forgot to give the bill and Neeraj does not make the payment by the due date and the bill is dishonored. Based on the provision of Negotiable Instrument Act, examine whether Nisha's presentment or presentation of the bill of exchange to Neeraj's assistants, is it valid or invalid? Of course, it is invalid, people. You have to give it to the person, that is drawee himself, or to any other person authorized by him. You cannot give it to any random person, even if that person is an assistant or anyone. If they are authorized to take it, you give it. If not, people, you cannot give it. And hence here, yes, not possible. Okay, explain circumstance. Bailment may be terminated. Concept of right of resale. Then easy one, Nothing complicated here. I hope it was easy and breezy. Okay. Next one. I hope you guys are able to answer the questions, da. Okay. Kashish was running a business of artificial jewelry since long. He sold his business to Naman. Kashish was running a business of artificial jewelry. He sold his business to Naman. Kashish sold his business to Naman. Okay. Naman made an agreement with Kashish not to carry on the business with artificial jewelry and real diamond jewelry in that area, and for a period Naman made an agreement with Kashish not to carry on the business of artificial jewelry and real diamond jewelry in that area, and for a period of next 1 year. After 2 months, Kashish opened a showroom for real diamond jewelry. Real diamond jewelry. Naman filed Naman filed a suit against Kashish for closing the business of real diamond business as it was against the agreement. Whether Kashish is liable to close his business of real diamond jewelry following the provisions of Indian Contract Act. Naman made an agreement with Kashish not to carry on the business of artificial jewelry and real diamond jewelry. Correct? Later on, what did he start? He started real diamond jewelry. Sir, whether the restriction was valid or invalid, restriction was reasonable. I cannot carry it in that area for 1 year. After that, can I carry? Yes, I can carry. Now, in this case, people, whether is the restriction valid or invalid? The restriction is valid. So, can this person can the person carry out? The answer is no, you cannot, because you have clearly agreed that you will not carry on this business of Naman made an agreement with Kashish not to carry on the business of artificial jewelry and real diamond jewelry. But there is only one thing here, people. I'll tell you both, reasonable and unreasonable. I am doing artificial jewelry. That is my business. Why am I stopping you from doing real diamond jewelry? Now that is an unreasonable ground. I can stop you from doing something which I am doing. I can stop you. I can say don't do. But why am I telling you not to do something which is nowhere related to me also? That becomes unreasonable. So on this ground, I will say, people, yes, Kashish is liable to close his business. Whether Kashish is liable, the answer is no. Kashish is not liable because the real diamond jewelry is nowhere in competing business. So the restrictions in that, people, is invalid. Clear? Good question. Okay. Albert obtained 2 loans of 3 lakh and 4 lakh respectively from a reputed bank. Out of these 2 loans, a loan of 3 lakh was guaranteed by Robert. Okay. There were 2 loans taken in since. One is 3, one is 4. Okay. And in this 3 lakh loan was guaranteed by Robert. Albert sent 2 lakh to bank but did not intimate as to how this amount to be paid. So I have repaid 2 lakh, it seems. I did not tell to which transaction to be taken. People, appropriation of payment, people. First, it will always be the choice of the debtor. If debtor is silent, then go as per the circumstance. One is 4, one is 3. So there is nothing for circumstance. The third one is, people, when the debtor is silent, people, the creditor can choose any order of payment. It is his choice. Even if creditor is silent, people, always go in FIFO. That is first in, first out. Okay, the bank appropriated the whole of the money towards 4 lakh. The bank took it towards 4 lakh, it seems. Why? Of course, because for 3 lakh they have guarantee. For 4 lakh they don't have guarantee. So he argued with bank that repayment amount should be first adjusted towards the guaranteed loan. That is, he's telling, no, what it is right, what it is wrong. You have to first set off the money towards 3 lakh and not towards 4 lakh. Now the question is, people, whatever is contention, is it valid or invalid? Of course, invalid, people. When you were silent, when you repaid the loan, that person, the creditor can set it off against any order of his choice. So your contention will be invalid. Next one, Parasnath Infra Height Limited is a public company and having 215 members, which 20 members were employees. Okay, 215 members. Limited means it's a public company. 20 members are employees. Were employees in the company during, when were the employees? From 1st June 2022 till 30th June 2024. Only during this period they were employees, it seems. They were allotted shares in Prashant Infra Limited on 1st April 2018. See here, they were employees from 2022 till 2024. But when did they become shareholders? They became shareholders even before they were employees. So I think they will ask you people, can a public company get converted to a private company? They have 215 members. Is it possible? In 215, 20 members are employees. Possible? That is what they would have asked you. Which are held by them today, that is 31st August 2024. Now the company wants to convert itself into a private company. State with reasons whether Prashant is required to reduce the number of members under the provisions of Companies Act. Is it required, people? The answer is it required? Answer is yes, required. Because they became a shareholders of the company even before they were employees. So under private company definition, who are excluded? The employees who are also the members of the company. So people, in our case, the employees got the shares even before they were employees. So can I exclude them? Answer is no. Can I include them in the count of members? Answer is yes. So 215 will be considered as 215 only. Done. Okay. Priyansh ordered 600 tins of apple juice from an American company, Am Juice Limited. The company informed that the tins would be packed in the boxes, each containing 50 tins. Company informed that they will pack it in each containing. Okay. On delivery, it was found that a substantial part was in boxes containing only 30 tins. They said we will pack in 50, but they have packed 30. Priyansh rejected the whole order as the tins were not packed according to the description. Okay. State with reasons whether Priyansh can avoid the contract under Sale of Goods Act. Possible? Yes, possible. Because you have given the description that I'll be selling it in the pack of 50, you have sold it in the pack of 30. So can I reject? Yes, people. Possible, provided that was agreed between the parties. That is 50-30. So is it possible? Answer is yes, possible. Both LLP, okay. Rahul and Kapil are partners in Measure Saxena Marble House. Rahul purchased 100 shares of reputed company in his name, but he made the payment from firm's account. One of the partner purchased the shares, it seems. He took the shares, but the money was paid from the partnership firm's account. Rahul did not consent to Kapil before acquiring the shares, referring to the provision of Indian Contract Act. Whether shares purchased by Rahul constitute a property of the firm? Answer is yes. What would be your answer if Rahul debits himself in the accounts books of firm and become a debtor of the firm? Meaning, if I'm, instead of the firm paying, I will say, I will only pay money. Give me some time. If it is shown as a debtor, people, then of course it is a valid contract, then no problem. The next one, Suraj Pharma Limited, a public company, its articles of association empowers the managing agents to borrow both short-term and long-term loans on behalf of the company. Mr. Smith, the director of the company, approached Easy Finance Limited, a NBFC, for a loan of 25 lakh in the name of the company. The lender agreed and provided the above said loan. Later on, Suraj Pharma Limited refuses to pay the money borrowed on the pretext that no resolution authorizing such loan have been actually passed by the company, and the lender should have inquired about the same prior to the providing of such loan. People, if you remember, people, doctrine of indoor management, we need not have to check whether the management procedures are done by the company or not. If you guys remember the case law also, people, Royal British Bank versus Turkyan's rule. Can the company reject its claim? Answer is no. Because if you have clearly written in AOA, this is my limit, then it will be binding. If you have not mentioned the limit at all in AOA, then how will the person who is an outsider, how will he know about the restriction? Agreed? Okay. XYZ was incorporated to hold the patent for a new product. Patent means dormant company. Okay. The company is expecting to start its commercial production within the next 2 years. In the meanwhile, for timely installation, the company has placed the purchase order for plant and machinery with a down payment of 1 crore. Possible, significant accounting transaction. Referring to the provisions, whether the company can go for acquiring the status of dormant company, of course no. Because people, significant accounting transaction. So it is not an inactive company. So a company cannot apply for dormant status. Nitin appointed Shiv as his agent to transport apples from Shimla to Delhi. Due to heavy rain in Shimla, Shiv was stranded for more than 7 days. Shiv was not in position to contact with Nitin. To save Nitin from loss, Shiv sold all the apples in the nearby market below the market rate. Explain with reference to Indian Contract Act, can Nitin recover the loss from Shiv? Not possible, people. Agency by necessity. If at all the agent is not in a position to speak with the principal, and if the agent has resorted to the best possible alternative action, whatever the agent does, people, principal will be liable. So principal cannot recover the loss from the agent. Agent by necessity. Explain the concept for presentment. What do you understand by law? Okay. Mr. Shankar sold 1000 kgs wheat to Mr. Ganesh on credit of 3 months. Wheat was to be delivered after 10 days of contract. After 5 days of a contract, a friend of Mr. Shankar secretly informed him that Mr. Ganesh may default in payment. See, it is to mislead you. On the information of friend, Mr. Shankar applied the lien and withheld the delivery. Referring to the provisions, state whether Mr. Shankar was right in his decision. Was he right? Answer is no. When can you exercise right to lien? Whenever the goods are sold on cash basis, whenever the goods are sold on credit basis, but the period of credit is over, whenever the person becomes insolvent. First one, people, it is not sold on cash. So first scenario is not. Second one, it is sold on credit 10 days and you are doing it within 5 days only. So the credit period is not yet over. And people, the friend has said he may default in payment. That means they have not used the word insolvent and the word is may. So you are not sure yet. So because of these things, people, so whether Mr. Shankar was right in decision, answer is no. What would your answer be? See, if he became an insolvent, then yes, you can invoke the right of lien. Clear? Done. Partner in a firm may be classified into dormant partner, nominal partner in profits or holding out. Okay. Sachin bought 1000 kgs sugar from Saurabh for 40,000 on 3 months credit. For this purpose, Sachin issued a promissory note to Saurabh on the same date, payable after 3 months. On the date of maturity, the promissory note was dishonored by Sachin. Saurabh filed suit for the recovery of the amount plus fees of advocate paid by him. Referring to the provision of negotiable instrument, what amount could be recovered from Saurabh from Sachin? Of course, people, you can recover 40,000. That is the amount mentioned on the bill. You can also recover advocate charges, court fees. All of this can be recovered. Yes, possible. The third thing, you are also entitled to an interest at the rate of 18% per annum. Because if you had given me money today, it will be 1 crore. If you are giving it to me after 1 year, I would have utilized it for some other purpose. I would have invested in my FD. I would have got at least some rate of interest, no? Hitting it up. Okay, explain the done. Clear? I hope it is easy and understandable. Nothing, no complicated question as such spotted yet. Mr. A was running an orphanage. His friend Mr. S, a philanthropist, agreed to donate rupees 2 lakh for treatment of a child who was suffering from cancer. On emergency, Mr. A incurred 1.5 lakh on treatment of child. Now Mr. S refused to pay Whether Mr. A can claim 1.5 lakh from Mr. S possible? Case law, which case law? Kedarnath versus Gori Mohammed. So people, if you remember, what is this coming under? Exceptions to quid pro quo. Charity. So will charity become a legal obligation on you? Answer is yes, charity is a legal obligation provided the other party has undertaken some liability. Based upon your word, if the other party has undertaken some liability, it becomes a debt you have to pay. Mr. L let out his residential house to Mr. M for 50,000 per month for a period of 1 year. According to the rental agreement, electricity bill will be paid by Mr. L. But Mr. L could not pay electricity dues up to 5 months due to his financial hardships. The electricity board sent the notice of disconnection. If it is not paid within a week's time, to avoid all this, Mr. M paid the electricity bill of 50,000 with penalty. Later on, L refused to reimburse 50,000 and argued that he has paid bill voluntarily because of his own interest. Decide with the reference to the provision of Indian Contract Act. People, they have made your life very easy. Payment made by an interested person. That's the provision. If the landowner does not pay, they will they will seize that particular property, or they will remove the fuse, because of that even the tenant also is suffering some loss. In that case, don't you think I will suffer some loss? So to avoid that, if I am making the payment, of course people, I can recover the money from you. So will I be able to recover? Yes, payment made by a interested person. Quasi contracts, yes or no? Okay. XYZ Limited was incorporated to hold the patent for a new product. Company is expecting macha cut copy paste, same thing, dormant company, plant and machinery, 1 crore, cannot be considered as a dormant company. Mike LLC incorporated in Singapore, having an office in Pune, India. Analyze whether Mike LLC could be called a foreign company. What is a foreign company? A company which is registered outside India, a body corporate which is registered outside India, which has a place of business in India and conducts any business activity in India, it will be considered as a foreign company. And hence Mike LLC is a foreign company because it is registered outside India. It has a place of business in India. It is a foreign company. State the modes by which a partner may transfer his interest in the firm in favor of another person. Okay. Sony, a friend of Priya, wanted to buy her two-wheeler. Priya agreed to sell her two-wheeler to Sony, and it was decided that the price of her two-wheeler will be fixed by Priya's father, who is an auto dealer. Priya immediately handed over the keys to Sony. However, Priya's father refused to fix the price as he did not want Priya to sell her vehicle. Priya expressed her inability to sell the two-wheeler to Sony and asked for return, but Sony refused to return the same. Explain, can Priya take back the vehicle from Sony? Will your answer be different if Priya had not handed over the vehicle to Sony? People, this is nothing but people, ascertainment of a price. It will be first decided based upon the course of dealing between the parties, based upon the agreement, or based upon the third valuer or the third party valuation. So if a third party, we have said that he will give a value, based upon that we will enter into a contract. But remember people, if at all anyone does any activity because of which the third party is unable to do the valuation, in such case such contracts can be avoided. That is one, remember. Second one people, whenever the goods has been transferred, whenever the possession has been transferred, in such case people, the buyer is expected to pay a reasonable price. You cannot avoid the contract. So in this case, can Priya take back? Answer is no. They will pay a reasonable price. Will your answer be different if Priya had not handed over the vehicle? Yes, my answer will be different. In such case, the contract can be avoided. Clear? Done. LLP, okay. P, Q and R formed a partnership agreement to operate motor business along specified routes for a duration of 12 years. After operating the business for 4 years, it was observed that the business incurred losses each year. Despite this, P is determined to continue the business for the remaining period. Examine with reference to the Indian Partnership Act, can P insist to continue the business? If so, what options are available to Q and R who are reluctant to continue the operating business? First thing remember, can P continue the business? Answer is yes. Because it's for 12 years. Only 4 years have passed. So can we continue? Yes, as per the agreement, we can continue. Sir, if you do not want to continue, what is the alternative Q and R has? First thing, mutual agreement. All of you guys have to agree and mutually dissolve the firm. If not, people go under the court's route. Perpetual losses. One of the ground for dissolution. The court may order for dissolution order. A and B operate a textile merchant business in partnership. Mr. A finances the business and is a sleeping partner. In the regular course of business, B acquires certain fabric goods belonging to C. However, B is aware that these goods are stolen property. Despite this knowledge, B proceeds to purchase and sell some of these stolen goods. Moreover, B records the proceeds from these sales in the firm's books. Now, A wants to avoid the liability towards C on the ground of misconduct by B. In the light of provisions of the Indian Partnership Act, discuss the liability of A and B towards C. Always remember, people, any wrongful act done by a partner, all the partners will be liable. Partnership firm will be liable. Even though you are a sleeping partner, acting partner, it will not make any difference. In our case, even though you are a sleeping partner, this person's liability will continue. It will not come to an end. XYZ is a company incorporated under Companies Act 2013. The paid up capital is as under. Okay, XYZ Limited. Oh, they have not given anything. Okay, XYZ. In this, Government of India holds 20, plus Government of Tamil Nadu holds 10, 30. Rajasthan 10, 40. LIC don't count. This you don't count. As per above, whether XYZ Limited be called as a government company? Answer is no. People, what is a government company? Where central government or state government or state and central or state governments hold more than 51% of the total voting power, total paid up share capital. We call such company as government company. Nowhere it says you need to add these two in the definition. So total capital is 40% and on those grounds we can say it is not a government company. M and N holding 70 and 30% of shares in the company both die in an accident. Perpetual succession, people, same thing. The company will not come to an end. Company can still continue. Explain in brief with reference to the provision of Indian Contract Act. What are the rights? Okay. Mr. J entered into an agreement with Mr. S to purchase his house for 20 lakh. Within 3 months, he also paid 50,000 as token money. In the meanwhile, in an anti-encroachment drive of the local administration, Mr. S's house was demolished. When Mr. J was informed about the incident, he asked for the refund of token money. Referring to the relevant provisions of Indian Contract Act, state whether Mr. J is entitled to the refund of the money. People, they are asking you as per Indian Contract Act. Do not get confused between Sale of Goods Act, transfer of ownership. First thing, Sale of Goods Act can never have immovable property. They have clearly given you Indian Contract Act. Now, what has happened? Indian Contract Act, contract is entered, but the effect is in the future. So it's an executory contract. Now, people, after the contract is entered, something becomes impossible to perform. What will happen to the contract? Contract becomes void due to impossibility of performance. Why? Because of change in law. And in such case, what happens? It's a void contract and hence the contract comes to an end. Whenever a contract becomes void, remember, whatever advantage the parties have received, the parties are expected to return the advantage received. So you have received the token advance, the money will have to be received. You have to return the money. 50,000 will be given back. Rama directs Shams to sell laptops for him and agrees to give Sham 11% commission on the sale price fixed by the Brahma for each laptop. As Government of India puts restriction on the import of laptops, Rama thought that the price of laptops might go up in near future, and he revokes the Sham's authority for any further sale. Sham, before receiving the letter at his end, sold 5 laptops. When will agency come to an end? When it is communicated to the agent, or for the third party, when does it come to an end? When it is communicated to the third party. So here, before it is received, he reads about it, he gets to know about it. He has already sold 5 laptops. Sham asked for 11% commission of 5 laptops at 1 lakh each. So what will be my commission? Whether the sale of laptops after revoking Sham's authority is binding on Rama. So people, after it is communicated, people, after you are aware of it, then people know you cannot bind. But after you are aware of it, will you be able to recover the commission? Yes, sir. How much, people? 5 laptops you have sold for 1 lakh rupees into your commission is what? 11%. 5 lakh into 11%, how much? 55,000. Correct, no? That will be my commission. Write down, see, calculate and show. Inchoate. Okay. Ram sells 200 bales of cloth to Sham and sends 100 bales by lorry and 100 bales by railway. Sham receives delivery of 100 bales sent by lorry, but before he receives the delivery of 100 bales sent by railway, he becomes bankrupt. Ram, being still unpaid, stops the goods in transit. The official receiver on Sham's insolvency claims that goods decide the case with reference to the provision of Sale of Goods Act. So people, there is one whole contract. In that 100 was sent by lorry, 100 by railway. Lorry has reached, railway has not reached. The person has become insolvent. Can I exercise my right to a stoppage in transit? Answer is yes. For the remaining goods in transit, I can exercise right in transit. Classify the following transaction according to the types of goods. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. So it is already selected and set aside. Ascertained goods, people, identified goods. Specific goods identified. A agrees to sell to B 1 pack of sugar out of the lot of 100 packets. Agrees, meaning in the future. So it is unascertained goods. Bulk. T agrees to sell to S all the apples which will be produced in his garden in the next year. That means, people, future goods. Referring to the provision of Negotiable Instrument Act, Aman drew the bill of exchange on Baban. Aman drew on Baban, who accepted it, and payable to Magan. Payable to Magan. Magan endorsed the bill to Gagan. Okay, Magan, what are they doing there? Gagan endorsed the bill to Akash. Abba. To be delivered. Okay, Gagan endorsed the bill to Akash to be delivered to him on the next day. Okay, Gagan endorsed, meaning he has signed. And the delivery is to happen tomorrow. However, on the death of Gagan on the same day, his only son Ankit delivered the bill to Akash. So Gagan did not deliver, Akash delivered. On presenting the bill on the due date, the Baban refused to pay, explaining the importance of delivery negotiation, decide whether Akash can enforce the payment of the bill of against Baban on the previous parties or not. Remember, people, endorsement is complete only after signing as well as transferring. Delivery of instrument has to take place by the party only. Upon the death, people, you just like that cannot give away the instrument. That cannot be considered as delivery. It is the same party who needs to give, not the one who has passed away. So no, it is not valid. Understood? Reliable Limited, an Indian company, is a global leader in petrochemical products. For payment of the sale price of machinery imported from Alex Manufacturing Limited, a USA-based company, the Indian company drew a bill of exchange on Manish, a resident of Mumbai, who accepted the bill at Mumbai payable to the exporter in Los Angeles, USA. decide whether the bill of exchange is inland or foreign instrument. Whether it is an inland or foreign instrument, we had seen this in our revision on all the place, people. Inland and foreign instruments are important. First thing you guys have to see, people, whether the bill is drawn in India. It's an Indian company, so of course it is drawn in India. If that condition itself is not satisfied, then close your eyes and write off foreign instrument. Okay, next one. Next two conditions I have to see is what? If it is payable in India or if the drawee resides in India. So this is mandatory. In these two, any one has to be satisfied. So they're telling you drawee resides in India. So one condition satisfied, one condition satisfied. So two conditions satisfied. Hence it is a inland instrument. Done. J, a wholesaler of premium basmati rice, delivered on approval 100 bags of rice of 10 kg each to a local retailer on a sale or return basis within a month of delivery. The next day, the retailer sold 5 bags of rice to a regular customer. A week later, K informed the retailer that the quality of rice was not as per the price. The retailer now wants to return all the rice bags to J, including the 4 bags not used by K. Can the retailer do so? People, sale or return basis. When does the ownership pass? Whenever you signify your approval. Next one, people, you keep the goods beyond the returnable period. Third one, people, you do something equivalent to an acceptance. In this case, what happened? A has sold the goods to B on a return sale or return basis for a month, 1 month. Now B further has sold it to C. Now when can you further sell it to C, people? As per the third condition, when you think that product is yours. So he has sold 4. So out of 100 people, I can return 96, no doubt, but I cannot return these 4 because on that you have already exercised your ownership. So it is the ownership is already passed. That's all done. Next one. X was running a business of car on lease. One fine day, Y came to hire a car for 10 days for his business tour from Delhi to Amritsar. X offered him a Honda City for 50,000 for 10 days on a condition that petrol and toll expenses will be borne by him. Okay. During the journey, engine of car was choked. Y has to spend 10,000 rupees for repair of the engine. Extraordinary expenses, the bailier only has to pay. When he was coming back from Amritsar, the brakes of the car were not working and a major accident also happened. Y was admitted to hospital and paid a bill of 5 lakh rupees on recovery. Y asked X to compensate him the hospital charges for car and hospital expenses amounting to 60,000. So will you get it, people? Yes, you will get it. Extraordinary expenses, whenever the bailment is non-gratuitous bailment, meaning if the bailment is for hire, whatever are the defects, whether known or unknown, you will be liable for those defects. So can I recover? Yes. What and all I can recover? I can recover every extraordinary expense. Meaning here 10,000 is repair cost, I can recover. 50,000 hospital cost also you can recover. So yes, I can. Evergreen Private Limited has 9 directors on its board of directors. The company's articles of association currently state that the quorum for board meeting shall be 1/3. Same thing, people, which we already seen, entrenchment of articles, public company, special resolution, private company, 2/3. State with reasons whether the following companies can be treated as small company. STS Private Limited having a turnover of 10 crore and the paid up capital of 1 crore. Paid up capital is 1 crore. That is 1 lakh equity shares. Out of these, 60,000 shares are held by UV. That means STS is a subsidiary company and hence it cannot be a small company. ZX Limited having a paid up of 3, turnover of 35. ZX Limited, see, name says limited, that means public company. A small company means a company other than public company. So no, it cannot become a small company. P sold certain antique items to Q for 3 lakh on 13th December 2024. As per the terms of agreement, 75% of the amount was to be paid within a week and balance 25% was to be paid till 31st December 2024. X appointed his agent R to take delivery of the goods after the payment of first installment. Q transferred a sum of 2,80,000 in the account of P through NEFT on 18th December 2024. Balance has to be paid within 31st December. Okay. Which was credited in P's account on the same date. R failed to take the delivery of antique items due to medical emergency. By the meantime, Q failed to make the payment of the second installment till 31st December. On 10th January, Q's agent came to take the delivery of the goods, but P refused to give. Can I exercise the right to lien on 20,000 rupees? Is it possible? Of course, I can exercise, people. The due date is 31st December. Now the date is 10th of January. Can I exercise? Of course, I can exercise because the credit period is over. Right to lien can be exercised, valid. An auction takes place in Delhi for antique items. It is notified to the bidders that the sale will be completed only when the hammer of the auctioneer hits the table and he announces you are the highest bidder. During the auction, L bids for an antique sculpture worth 8 lakh. The hammer falls, but announcement cannot be made as the auction suddenly stops before the auctioneer can utter any word. It is notified to everyone that there has been an unexpected rise in the market price of the particular sculpture and therefore it will not be sold on the particular day. L contends that the auctioneer is bound to sell the sculpture to him at the price he bid because once he bid the highest price, the auction and the hammer fell, the auction sale was complete. Auction sale will be complete, people, based upon the customary actions that the person has followed or any other means. So in case it is clearly written, people, 3 times of hammer and you are the highest bidder had to be announced. It is not yet announced. And hence, people, the sale is not yet complete because it is not yet announced, which is customary. Simple. PQR are partners in a construction of PQ. P buys cement. Same thing. We need not do it again. The object clause of MOA authorized the company to carry on the business of trading in property in Gurgaon. Since the company was not doing well, the directors of the company in recent board meeting planned to diversify the business and enter into a construction business. For this, they borrowed a sum of 5 crore from Magnum Finance for the members of the company. Company refused to repay the loan. According to the problem, what is the recourse available to Magnum Finance? Okay. People, yes, it is ultra vires transaction. If you have borrowed the money for any other purpose, it is the ultra vires transaction. Company will not be liable. However, if company has taken the benefit of the money so borrowed, meaning we have borrowed 5 crore, in that some 2 crore rupees was taken a benefit by the company to repay some other debt. In such case, people, my liability will not come to an end. My liability will continue. So I will have to repay in such cases. Though it is ultra vires transaction because the company has taken the benefit here. S&M Limited was registered in 2021 with share capital 50 lakh divided into 5 lakh. Section 8 company promoting, okay. Company earned huge profits. Demanded for dividend, people. Possible, definitely not possible. Okay. Okay, explain the validity of the following agreements. Marriage Bureau, which we already seen. Bharat agrees. White Bull, which was dead. Mutual mistake, we have seen. Rishabh sells the goodwill. Omkar, which we have seen. Local limits, valid. A property worth 2 lakh was agreed to be sold for 25 on unsound mind. We have seen. Done. MNO Limited, a supplier of electronic components, entered into a contract on August 1st, 2023 with PQR Limited for sale of thousands units of microchips. Microchips, people, already done. Correct, huh? Okay, A purchases a motorcycle from B and uses it for some time. It turns out that motorcycle sold by B to A was stolen. What will you do, da? I need to return the goods. I need to take back the money. Implied condition as to the title. Classify the negotiable instruments. A promissory note made in Kolkata, payable in Mumbai, inland only. Two conditions. Where it is made, payable, and where does a drawee reside. Made in Varanasi, on a person resident in Jodhpur, drawee resides in India. Yes, people, it is inland. Agra draws a bill of exchange in Agra. Residing in also Agra, bills of exchange also drawn in Agra only. A promissory note is made in New York, drawn outside India by a resident of New York. Two conditions also not satisfied. So I'll call it as foreign instrument. A bill of exchange is drawn in London on a person residing in Dubai. So two conditions not satisfied. Foreign. Done. Classify the following transaction according to the type of goods. A wholesaler, 100 bale, agrees to sell ascertained goods, existing goods. A agrees to sell 1 packet of sugar, unascertained goods. Done. The last one, sir. Rahul owns an electronic store. Pankaj visited the store to buy a water purifier priced at 54,000. He specifically requested Rahul for a purifier with a copper filter. As Pankaj wanted to buy the purifier on credit with the intention of paying in 9 monthly installments, Rahul demands a guarantor for the transaction. Suraj, a friend of Pankaj, came forward and gave the guarantee for payment of this water purifier. We'll see. Suraj came forward and gave the guarantee for payment of water purifier. Rahul sold Pankaj a water purifier of a specific brand. Pankaj made payment for 4 monthly installments and after that became insolvent. Explain with reference to Indian Contract Act the liability of Suraj as a guarantor to pay the balance price. Of course, people, it was 54,000 rupees. He has paid 4 installments. Correct? How much is each installment? They have not given. Okay, he has agreed to pay 54,000 divided by 9. 9 installments. You see how much will come per installment. Yes, 9 5s are 45, 9 6 are 54. So you need to pay 6,000 rupees every month. He has paid 4 installments. So he has paid 24. That is remaining people how much? He has to pay 30,000. When the borrower fails to pay, the guarantor will have to pay 30,000. What will be your answer if Rahul sold the water purifier misrepresenting it as a copper filter? In such case, people, the liability of principal lender also will come to an end. Then the liability of the surety will also come to an end. A company DEF Limited as on 31st March 2024 had a paid up capital of 1 lakh. 10,000 shares. In June 2024, okay, once again. DEF. They have paid up capital of 1 lakh. Okay. They issued another additional shares of 1 lakh. So now it is 2 lakh. Out of 10,000 shares, 5,000 shares were issued to MNO Private Limited. Out of this, MNO Private Limited are holding how much? Total 5,000 shares. That is 50,000. MNO is a holding company of JKL. MNO is a holding company of JKL. Okay. Now JKL Private Limited claims the status of being a subsidiary of DEF Limited as being a subsidiary of its subsidiary MNO Private Limited. No, people, these are not subsidiary and holding. Nowhere they are related. Of course, they are not related. Okay, they are not related. No, it cannot be called a subsidiary company. State the relationship between DF and MNO. These two people. What is the relation? Who can tell? Of course, the relationship between them is people, associate company, because they are holding 25% of shares in the DF Limited. What is an associate company? A company which holds in other company a significant influence. Now, what do you mean by significant influence? Significant influence means people, something which is at least 20% but not more than 50%. Ashish, a trader, delivered camera to Mohan, on sale or return basis. Ashish delivered a camera to Mohan on sale or return basis. Mohan delivers the camera to Raj for sale for cash only or return basis. Raj delivered it to Vikas on sale or return basis without paying cash to Mohan. So R has not paid cash to Mohan. This is not paid. The camera which was in possession of Vikas was lost. Vikas lost the camera. Left though he exercised due care, meaning what? He has taken proper care. If not, you can say V is responsible. Referring to the provision of Sale of Goods Act, analyze the situation, advise whether Mohan, Raj or Vikas are jointly or severally liable. Who will be liable? People, Ashish gave his camera on to Mohan on sale or return. On sale or return, when will the ownership pass? Whenever you accept, whenever you keep the goods beyond the period. The third one, people, you do something equivalent to an acceptance. Here you have done something equivalent to an acceptance. You will further sell it only when it is yours, right? Yes or no? So here, sir, he has further sold it to Mohan. So, sir, ownership is transferred to Mohan. Agreed? Okay. Now Mohan is the owner. Now Mohan has given it to Raj, but Raj has not paid the cash. So there is a clear condition. Until the condition is not met, right of disposal is reserved. So ownership is not yet transferred. Money is not yet paid. So people, definitely Raj did not become the owner. So did Vikas did not become the owner. So whose responsibility it is ultimately? The entire responsibility is on the Mohan. Rest of them are not liable. Akash of Jaipur sold 100 smart TVs at 50,000 per set to Barun. He delivered the TV sets to Chirag, a transport carrier, for transmission to Barun. Barun further sold these 100 TV sets to Sarthak. Akash sold to Barun. Okay. Whenever names come in your exam, it is your responsibility to first write down it like this. And don't write on question paper. Take pencil and write it in your answer sheet only. After everything is done, erase. Okay. He delivered the TV sets to Chirag, a transporter. Okay. It is given to Chirag, a transport agent. Okay. Barun further sold this to Sarthak. Ababa. On reaching the goods at the destination, Barun demanded delivery, but Chirag wrongfully refused to deliver. People, simple da. See the words. This is what I call it as keywords. Whenever the goods are wrongfully refused to deliver by the carrier, the transit comes to an end. Agreed? That is why he failed to deliver the TV sets to Sarthak and suffered a huge loss on account of non-delivery. Akash came to know about this. He directed Chirag to stop the delivery to Barun and re-deliver the goods to him at Jaipur. Answer the following. Whether Akash has the right to stop the goods in transit? No. Transit has come to an end. Whether Barun can claim loss? Answer is yes, Barun can claim loss. Possible. Ram wants to incorporate a company. Okay, how you follow, you file form spies and all. Okay, done. Okay, Ram and Sham are partners in a partnership firm, RS & Co. Gaurav, a renowned businessman, is their common friend. Ram and Sham are the partners. Gaurav is their common friend. Okay. Ram introduced Gaurav to Sahil. Ram introduced Gaurav to another person called Sahil, a supplier, as his newly joined partner. Gaurav, knowing that he is not a partner, preferred to keep quiet. What do you mean by it? What is the answer? Partner by holding out. This information about Gaurav being a partner of the firm was shared by Sahil with another businessman. Sahil also told it to another businessman, it seems. Who? Madhav. Sahil told Madhav that, hey, you know what? Gaurav is their new partner. Who told? Sahil told. Next day, Sahil supplied the raw material on credit and Madhav lent 5 lakh to the firm for a short-term period. So now what happens? Sahil and Madhav both have done a contract with RS. So the question is, people, simple. So if something happens, is Gaurav responsible for this contract? If yes, to whom is he responsible? Sahil or Madhav also? Of course, people, wherever he had an opportunity to deny, only with them he will be personally liable, not to the party whom they have further communicated. For Madhav, I will not be liable. For Sahil, I will be liable. Because with Madhav, I did not behave anything. Sahil was the person who told, not me. On admission as a new partner, Ashwin agreed to be liable for the existing debts of the firm by an agreement signed by all partners, including Ashwin. Examine whether Ashwin will be liable. Yes, people, you can be liable provided it's a novation. Only additional condition is that people, in addition to the partners, even the creditors also should agree to it, not only you guys. Here they have only said the partners will agree, and hence people know. This cannot be considered as a valid novation. MN Limited borrowed a secured loan of 5 crore from Star Bank to meet its working capital. Same thing, MOA, ultrawires. If you have used the money to repay, the utilization of the remaining 2 crore cannot be traced. The company's books of accounts show that the company has utilized a loan of 3 crore for repayment of its lawful debt. So even if it's an ultra-wires transaction, people, I can recover the money. Clear? After incorporation of Unique Private Limited on 15th May, the share certificates were issued to Arnav, Sohail and Suman, being subscribers to MOA of the company without affixing the common seal. Is common seal mandatory? Common seal is optional from 2015. In the place of common seal, who should sign? 2 directors have to sign. If a company has a company secretary, then 1 director and 1 company secretary have to sign. So without affixing common seal and under the signature of Arnav and Sohail, the directors of the company, Arnav and Sohail, so 2 directors, is it valid? Yes. The company has yet to appoint CS, so there is no CS. Is it valid? Yes, it is valid. What if a company has a CS? Then it will be 1 CS and 1 director. Mr. R extended a loan to Mr. D with XYZ as sureties. Each surety executed a bond with varying penalty amounts, X with a penalty of 10,000, Y with 20,000 and Z with 40,000. People, co-sureties. To what extent? People, okay, see, the total amount they have given is 70,000. But what is the total default made? 42,000. Remember people, as long as you can equally divide, you have to divide the loan equally. So 10,000, 20, 40 is the total difference, different amounts they have agreed. So to the extent of 10,000, all of them can be liable, correct? And there ends the first person's liability. Now still how much is pending? Still 12,000 is pending. Now the first person cannot be liable anymore. His liability comes to an end. The next person can be 20, 40. So I need to divide 12. So divide 12 equally. So what will be the liability? This person is 10k, this person is 16k, this person is 16k. Clear? Done. Important from exam point of view. Remember and go. X agrees to pay Y 1 lakh if Y kills Z. To pay Y, X borrows 1 lakh from W, who is also aware of the loan. So people, illegal agreements, agreements connected with illegal agreements will also be considered as void. So X agrees to pay Y 1 lakh if Y kills Z. So contract between X and Y directly it is illegal. X and W, because you are aware, W is aware that the money will be taken and given to this purpose. Any agreement connected people will also be considered as void. Karan agreed to sell his laptop to Vishal for a price to be fixed by Kiran, a hardware engineer. However, before the delivery, changes his mind and did not share any particulars and configuration of the laptop, which made her unable to do the valuation. So whenever any parties to the contract prevents the third party from doing the valuation, in such case you can avoid the contract, you can avoid it. You can also claim compensation. Vishal needed laptop for his project, so he promised Karan that if the laptop is delivered to him, he would pay a reasonable price for it. However, Karan decided not to sell his laptop to Vishal. Now Vishal wants to know from you, being a legal expert, whether Karan is bound to by his promise as he agreed earlier to deliver his shop. So people, if the possession is not transferred, people, then no, I need not have to pay the reasonable price.
If the possession is transferred, I need to pay the reasonable price. Miss Meenu went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price the same as 125 rupees per kg, to which she agreed. Miss Meenu insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon such a purchase. Controversial question. The shopkeeper showed her a bowl of rice as a sample. The sample exactly corresponded to the entire lot. Corresponded to the lot. Miss Meenu examined the sample casually without noticing the fact that even though sample was that of basmati rice, but it contained a mix of long and short grain. Now people, the cook on opening the bag complains, okay, now Miss Meenu wants to file a suit for fraud against the seller, alleging him of selling a mix of goods, cheap quality rice. Decide the fate of the case and options open to Miss Meenu for grievance redressal. Now why I am telling you controversial is people, in this MTP, which is in Jan series, they have said people it was Meenu's responsibility to check it properly, and because the sample corresponded to the bulk, Meenu will not get back her money. But if you go back any time before Jan, they have asked the same question in the exam also, they have asked the same question in the RTPs also, but the answer has been different. Why? Whenever you are selling the rice as basmati, there is a description and there is also sample. The institute itself in the past has given this particular question as sale by sample and description. The description is to be met. So when you say basmati, basmati has to be long grain rice. The institute itself had given. In this people, they have given a different answer. They have just referred it to sample and they have answered it. According to me, this question is wrong. The interpretation they have taken is wrong. Clear? Mr. Y issued a check for 10,000 to Mr. Z, which was dishonored by the bank because Y did not have enough funds in his account and has no authority to overdraw. Examine as per the provisions of negotiable instruments whether Mr. Y is liable for dishonor of a check. If yes, what are the consequences for such offense? 2 years of imprisonment or twice the amount of the check. This or that or both. Check is 10,000. So it can be 20,000, up to 20,000. What would be your answer if Y issued a check as donation? Remember, check bounce case can come only and only in the case of legally enforceable debt. Donation, no, gift, all this are not the valid grounds for, it's not the valid grounds for dishonor of a check. I cannot take it. Yes, sir. That's all, people. A quick revision of I don't know how many questions, but I hope, see, that's why I say seeing the questions will give you different perspectives of reading the same topic. Now, you might have read the same topic, but you might have read it in a different way. That's why I always say read multiple questions. So that's it for today. Tomorrow, let us meet again, people, with RTPs. Let us revise quickly 5 RTPs. And the last day, make sure you take, you guys are looking at and you guys are, learning something out of it. We will be practicing on how to write your answers. So thank you so much all. See you. Bye-bye. Okay. Now people, what is that? So today what are we doing there? What is that? Paper presentation. So we are going to have writing practice. So I should also write. Okay, let us write. Let us see how to present the answer. I'll try to present it the way that we are going to do now. In the exam, what are the key preferences that I'll be giving for a particular answer? And how do I make sure that the valuer sees these words specifically? And what is that I need to make sure I have to write? And what is it I can write in my own words? So what is that I have to take it from the book? What is it? It can be in my own words. That interpretation we'll try to see today. Clear? So randomly I asked the team to give me 3 questions. So we have taken 3 questions. Clear all of you? Okay, done. So we'll see in 3 questions how to write. And before even we see that, I'll tell you what are the certain mistakes that people will do, certain mistakes that you should not do. Always remember, people that end up in 195, 190, 192, the biggest problem in their life would be they have not taken the MCQs properly. Whatever is the risk you guys want to take, whatever ChatGPT has told you till now, risk is everything, whatever quotations you have seen till now, everything should go for MCQ. Your targets for MCQ should be, at least I'm telling you, is you have to score 60. I'm not saying you have to attend 60. You have to score 60. The moment you're getting 120 in your MCQs, people, the rest of the 2 papers where most of the people find it challenging, all that you need to get is 80, which is manageable. 40 to 45 is literally manageable, not even a competitive spirit at all. 40 to 45, easily manageable. But where will the problem come is, always remember, when you try to play the game equally, what will you do? Sir, it's okay even if I get in MCQ, if I get 40s also it's okay, 45 is also okay. Now you have a pressure to earn that marks somewhere else. Now where will you earn it from? So it has to be spread across. Your risk has to be spread across MCQ papers. That has to count. Risk it, take it, it's okay. We don't have a choice. Is this clear, all of you? That is the first thing. And second thing, you guys have to attend for all 100 marks. Sir, now law, I'm telling you, now you guys have started writing the tests. Correct? What is the number you guys are able to touch? You guys are writing 100 marks test whenever you are writing. Okay, how much you are able to complete? How many of you have actually written 100 properly? That is, I have written 100 marks. How many of you are able to write? This is the second thing I'm telling you. Writing 100, not scaring you. Writing 100 will sound like impossible. We can't touch 100 marks unless and until you guys have writing practice. So for people who are watching also, make sure you guys write at least 1 paper. Reality check. Your preparations are done by now. Now take a clock. Keep it in front of you. See how much time you guys are consuming to write 1 paper. You have to touch 100. Now if I say 100, you might touch 95. You might touch 90. Anyone who is going 80 or less than 80, no, pull up your socks. Then something fundamentally is going wrong. Then if you are getting 40, you're getting 40 on what? You're getting 40 not on 100. You're getting 40 on 80 because you wrote 80. So try to increase your speed. And how do we do that? Have targets. Have a clock. Have a target. First 1 hour, you guys have to write 30. Next second hour, you guys have to reach 30. The God has given you very special abilities. In the last 1 hour, you guys can write 40. In fact, you will write 50 also. But that last answer is prescription. That you only can read. She says, I also can't read, sir. Simply for sake of it, I'll write it. Agree, that is a reality. Now that's what we all do. Now how do you expect magic to happen? 80 cannot work. And this is what is the strategy. If you don't know, go to the next answer. Leave the page, go. Leave the page, go. And always remember, the first question should be the most confident question. Is this clear? And never write lengthy paragraphs. I'll be seeing few people writing lengthy paragraphs. Avoid that habit. Never write lengthy paragraphs. Who has patience to read all that? And remember, yours is not the only paper that person is going to evaluate. Let us show some consideration to them also. They are also humans, doing the same paper again and again. And you also know you can't read your handwriting. And you get offended. Hey, it's a reality. We know what our handwriting is. Yes or no? Put little effort. Instead of making your first handwriting look like, oh wow, and last handwriting will be amoebas. It's okay to have from the first question, have a normal handwriting, normal, legible. And wherever important, underline. Yesterday also someone was asking me, law, sir, should we quote sections? If you know, please quote. Please write. If you don't know, don't write. It's okay. I think I would have given you all that important section list. You guys got that? I think I'd given no. The app it's there. But all of you don't have. So you guys are all not friends now. Big boss. I got it. I'll only have it.
I got it for Mayadam itself.
So that is there. Then why all these things? Do little research. Important sections. I'm telling you, at least 40 to 50 marks that sections will come. How many of you have watched that most important topics? I'd done a video recently. All of you have watched? Illa, we won't. Yes or no? Yes or no, da? No, we won't. Watched Instagram yesterday. Watched Baba Banduru reel? You watched or not? Baba Banduru reel? Yes sir, that and all we should watch, of course. What sir, you and... Correct, I'm sorry. Hey, then why I am going and screaming there? It's for you only. Yes or no? See, when students are there, no, I will do all this. That's why I say I'll only do it with camera. They want content, let them take content. If not, all this will come. Simply somewhere the teacher will get a yo papa and all. That's where I'll start telling what is happening, what is going wrong. So start making utilization of all those resources. Some based on some scientific analysis, I said these can be the probable questions. Meaning I'm telling you what are the probable topics. Last second, don't leave them. Especially those people who say that, sir, I have left Indian Contract Act, it is okay. Is it okay, you will ask. Sir, I have left this chapter, it's okay. That is what the questions you will be asking. So at least in that case, see these topics and go. Don't leave those topics. Agreed? All of you? So make sure you do that. And whenever it's a direct question, never write in a big paragraph. Split it into points and write. Are you getting? And what is the format we follow? We always follow one format. Now let us imagine if we are writing indirect question. That is case-based question. What is the format we follow generally? We always follow. The first paragraph will be the opening statement. Will always be provision. Meaning whatever is the scenario they have given. In my first paragraph, I should not use any words, any names, nothing given in the question. Whatever for that topic. What does your book say? Cut, copy, paste you have to write here. Whatever your book says. My first paragraph will be that. My second paragraph will be facts. Facts is nothing but a synopsis of the question. What is that they are asking? Facts is nothing but summary of the question only. So your fact should always be short. Don't keep it lengthy. The last part is people, of course, there can be a scenario where some real life cases can be relevant for that particular question. In that case, you can feel free to write here, referring to the judgment that is given in case law. Which case law? You can refer that. The last part will be people conclusion. So this will be the format we will follow. The provision will be people, what is the law saying in my book? Cut, copy, paste. The next one will be people facts. That is nothing but the summary of your question only. The third one is if at all your question is relevant to any case law, write the case law. The fourth one is people conclusion. Conclusion is nothing but yes or no. Whatever they have asked you in the question, take that only and write. Keeping this in mind, let us answer 3 questions today. You guys also write, I will also write. Clear all of you? Hello? After the session is done, if anyone wants to show it, you show it, I can guide you. If not also, I'll be writing it here only. You can compare. Clear? All of you? Okay, let us write. Okay. Paridhi, a minor falsely representing her age. See, they have taken from RTP. Correct? This question has been there. You guys have already written. Okay. Paridhi, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Mittal, owner of MP laptops, for purchase of laptop on credit amounting to 60,000 on 1st August 2022. She promised to pay back the outstanding amount with interest at 16% per annum by 31st July 2023. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Paridhi was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she is a minor and now he can't recover even a single penny from her. She will be a major on 1st Jan 2025 and only after that agreement can be ratified. Explain by which of the following ways Mr. Mittal will succeed in recovering the outstanding amount with reference to Indian Contract Act. By filing a case against Paridhi, a minor, for recovery of outstanding amount with interest. By filing a case against Mr. Ram, father of Paridhi, for recovering of outstanding amount. By filing a case against Paridhi, a minor, for recovery of outstanding amount after she attains majority. That's the question. You guys also write, I will also write. Simultaneously will write. You don't copy, I will not copy yours. Don't do group discussion. Now write whatever you understood. Done? Meaning facts are registered? Yes? Okay. Or once you are done, we'll write simultaneously. Okay. All of you are able to write? Easiest question. No group discussion. Yeah. Whatever you think is right, write down. Done. 2 more minutes. Last minute, 1 minute. Done. The best part about ICU is that when you guys pass, the pass percentage will be very good. So in your next level of CA, you will have a very good group with you. So now exactly what happened previously for CA Foundation to CA Inter. A group of 8 people together will pass. So going to the next stage with a group is always the best thing. Okay, done now? Okay, so people, yes, what is your answers? How will I write? Now my answer will be people. First we should do like this. And then whatever we will write. Om and all. Correct? So after writing all that, they are not supposed to write all that. So coming to the answer, I'll write. So I can start the answer in any way. So how I'll start saying that as per section, which section? Section 11. If I know, I'll be writing section 11 of Indian Contract Act. As per section 11 of Indian Contract Act 1872, an agreement entered with a minor shall be considered as void ab initio, which means invalid from the beginning. Which means invalid from the beginning. Now I can write the answer in 2 ways. First, I can write off provision here only. I am giving you alternate number 1. What is my alternate number 1? And I'll write accordingly, the agreement with a minor shall have following rules. Following rules. And what is that? Rule number 1. What is that, people? A minor agreement. Now see what are the questions they have asked. Can I file a case for recovery of outstanding amount with interest? A minor is not liable for the agreements as such agreements are void. Correct? That's my first rule. Now what is my second question? See here. By filing a case against Mr. Ram, father, can a minor bind his guardian? I'll have to write that rule, and I'll be writing a minor cannot bind his guardians personally unless they have authorized in the capacity of an agent. Correct? That is, what if parents only have authorized the child as their agent? Can they do it? Can a minor become an agent? Possible? Possible. So what if a principal, that is parent itself, has appointed minor as an agent? Possible. In that case you can bind. So I cannot write it, you cannot bind at all. Okay, my third thing, what are they asking? By filing a case against Paridhi, a minor, for recovery of outstanding amount after she attains majority. Can I recover money after you attain majority? What is the word? A minor agreement can never be ratified. A minor agreement can never be ratified. So this is my provision. My provision and done. Hello. So cannot be. Can never be written. Oh my God. Oh, you said, sir, why did you write can be? I'm so sorry. I wrote can never be. Okay. So now I'll write, people. Now what are the questions? 3 questions they have. Now what is that? She'll be a minor, can be ratified. Explain by which of the following ways Mr. Mittal will succeed in recovering the outstanding amount. Now people, answering the question referring to the above provision, answering to the question referring to the above provision, the liability of Paridhi, Paridhi only, no, is as given under. Now what I will write? I will write my first scenario. They have given you no solution now. Conclusion 1. I will write what? By filing a case against Paridhi, a minor, for recovery of outstanding amount with interest. Can I recover? Answer is no. I'll write, people, Mr. Mittal will not succeed as agreement is void, and hence Paridhi is not liable to pay what they have asked, principal and interest. I'm so sorry, I just said principal. No shortcuts, so full form only you should write. Clear? My first solution is done. My second solution. What is my second solution? By filing a case against Mr. Ram, father of Paridhi, for recovery of outstanding amount, I'll write Mr. Mittal cannot recover any sum from the father of Paridhi as minor cannot bind guardians. Hello? What is the third one? Paridhi shall not be liable even after attaining majority as minor agreements cannot be ratified. Now my answer presentation is done. Now what I'll go back, I'll go and revisit. First thing I will always see, I will see whether have I missed answering any question. Because they have clearly given as serial number, the chances are that you will not miss the particular serial number, so you are always safe. But what if it is not in serial number? If it is in a paragraph, there are chances that you will always miss a part of a question. Go and see it once, especially the last 3 lines. See. Okay, now I'll come back and see, okay, everything done. Section 11, I'm confident about my section. I will underline. Now, is it a science? Is it Greek and Latin? I know what is important. Void ab initio. What do you mean by that? Invalid from the beginning. Underline. Okay. A minor is not liable for agreements. Such agreements are void. Agreement. Underline. Minor cannot bind guardians. Underline. Minor can never. Minor agreement can never be ratified. Underline. Understood? Now go to conclusion. Mr. Mittal will not succeed. Mr. Mittal cannot recover. Paridhi shall not be liable. That's the answers. And that is my answer. On 5, you will pakka get 5. You write this, value will come and hug you. Understood? Pakka na, one way of writing. Do you want an alternative or is this good? This good? We can go with this. Right, sir? You said no, you will help her. Write and go. Okay. Or I will write, my first statement will be same. Section 11. As per Section 11 of Indian Contract Act, minor agreements are void ab initio. Done. Now I'll write people coming to the same thing. Whatever you wrote here, you write the same thing. Answering the questions referring to the above provision. So I'll write people, the first scenario. Explain the provision, write the conclusion. Explain the provision, write conclusion. So what did we write now here? Section 11, Indian Contract Act, minor agreements are void ab initio. I did not write anything else. Now what is the first one? A minor agreement is void. An agreement with the minor is void. That will be my provision. I will write it as a conclusion for one. I will directly write people, what is that? An agreement with minor is void ab initio and hence a minor cannot be held liable. Is this clear? It's my provision. Now, see, that's my provision. It's a conclusion. Hence, Mr. Paridhi, whatever his name. Mr. Mittal cannot recover the principal plus interest from Paridhi as agreement is void. That is my first answer. My second answer. What is the second answer? Second rule. A minor cannot bind the guardians. unless expressly provided or authorized, and write the solution. Hence, Parithi cannot bind his father, so Ram will not be liable. Mr. Mittal cannot recover any money from Ram. Third one. So what are the two ways of presentation? Always remember, when I think the topic is common, minor agreement, it's common, I will establish all my rules in my provision only. And conclusion, I will directly write applying the provision to the conclusion. I will directly apply it. And I will say yes possible, not possible, not possible. One way. The second way of interpreting it is write down which section and write the conclusion and write every rule and then what the conclusion says. Rule and conclusion. Rule and conclusion. Both are valid. Now if you ask me which is more impressive, the impressive one, nothing like that. Both are good only. If you ask me specifically what can give you more marks, second one can fetch you more marks because you are clearly writing for this conclusion, this is the answer. For this provision, this is the answer. So there are 3 points. I am writing that only. Specifically I am writing. So this will have more weightage. But nothing like, okay, if you write that you will not get, not like that. Both are valid only. But this is more precise and to the point. Clear? Hello? If you want, I told you the answer will have 4th paragraph. The 4th paragraph is, I can always give a reference to a landmark judgment, Mohiri Bibi versus Dharmodas Ghosh. I can also include, there is an established principle that was derived from the case law, Mohiri Bibi versus Dharmodas Ghosh, that an agreement with a minor is void. Hello? Now where will I write it? If you want, you can add it here only before you write it. Is this clear? There only you can add. You want? Clear? Have I written properly? I'll get marks. I can pass. Now if you write like this, you tell me, is it? Now do you think I refer to the book language? If you see, these are the keywords I tell you guys inside the class. Based on the keywords only I wrote. Where is the law now? Where is law? Now you compare. More than sufficient. You'll pakka pass. Pass Allah, you'll pakka touch 60. Pakka. Are you getting the point? But what is the problem? Ratification. Word has to come from you. Guardian. Word has to come from you. The keywords you guys have to remember. Are you getting it? Okay, this is clear? Okay, second one. Rohan found a valet in a restaurant. He inquired all the customers present there, but the true owner could not be found. Ababa, which one? Find out. He handed over the same to the manager of the restaurant to keep the valet till the true owner is found. After a week, Rohan went back to the restaurant to inquire about the valet. The manager refused to return it to Rohan, saying that it did not belong to him. In the light of Indian Contract Act, can Rohan recover the valet from the manager? Right. I can write off directly. Yes, sir. Why, sir? All this. Tell me, do we have any section? Okay, let us imagine we don't know section. Do we know section? Finder of lost goods. Remember section 71? No. Yes, all these are important. Hey, minor row, wager row, all these are important. Wager what? Section 30. So remember all that. It is important. Yes, wager. See, way. W. W da. How I remembered as a student. This is a coin. Can you say heads or tails? You can never predict it. So uncertain. Wager. W. 3. Wager. Every Killadi da. Okay, understood? Now people, now how will I write? Let us imagine, let us take both the ways. Of course, we will not know sections for every particular question. In such case, what we will do? We will write as per the relevant section. Sorry, we don't know section, no. As per the relevant provision of Indian Contract Act 1872. What is the question? What is the provision now? The finder of lost goods assumes a duty of, what will be the duty of finder of lost goods? To keep it enjoyed. Then until that time, where should I keep it? Safe. So what is it called as? The finder of lost goods assume a duty of, what will be his duty? That one word, whoever tells it, I'll give you one chocolate. Eclair's chocolate, 1 rupee. Now I got your wallet. Your wallet I got. What will be my duty?
Assume it as your own. As your own.
Understood? Demand and supply. Demand is provision. Exact word. What we write, you understood? We will write, we put our name only, sir, there. So I'll be writing, as per Indian Contract Act, the finder of lost goods assume a duty of the bailee. That means what? Hence, the person who finds the lost goods will have the following responsibility. What is that? To take care of the goods. As or with ordinary prudence. Or you can say without negligence, with due care. You can write that point. Next one. Retain the goods until the true owner now, you know what I'm establishing? My second point I'm establishing, what is the point as per which I'm telling the cashier can keep the, sorry, who is that? The person who found it. As per which point I'm telling you can keep the goods. There has to be a point in the law, no? In minor you said, minor agreements cannot be ratified. As per that I am telling you, even after I become a major, I will not be liable. And I established a principle that minor cannot bind guardian. And that is what I am telling you, Ram will not be liable. So here, as per which rule you are telling, whoever finds it will be the true owner. This is the rule. Until the true owner is found, you can keep the goods with you. Whoever found it. That's what the rule is saying. So as per this I will write. Now what? You can go and answer. Should I? Provision is clear. Okay. Now I'll write people. Do we have any case law now? Do you have a case law? Which case law? Very good. Referring to a decided case law which shares similar facts. That is, which one? Holland versus Howler. Correct? Yes, sir. So, now this becomes my provision, my what is that? Referring to judgment, case law I have given. Now I'll write my conclusion. What is that? Referring to a decided case law. Now people, as per the provision as per the provision and decided case law, it can be concluded that now what I need to write in my summary, don't use your brain, copy paste what they have given. The manager refused to return it to Rohan, saying that it did not belong to him. In the light of Indian Contract Act, can Rohan recover the wallet from the manager? Can he recover? I will write concluded that Mr. Rohan can recover the wallet from the manager. And we remember in the class, if you guys see, after paying any lawful expenses incurred by the clear. This is my conclusion. This is my answer. Clear? Isn't it simple? Yes. Now go back again. Same duty. What? Do I know section? Underline. I don't know section. It's okay. But I have to establish. What is it? It is a rule of finder of lost goods. And it is a duty of a daily. Retain the goods until the true owner is found. Conclusion. Can recover. And remember, conclusion should not be your own words. Go copy paste. Every question will have the conclusion. Write it only. Can or cannot. Yes or no. And rewrite the same phrase. That's all done. Hello. Pakka. Okay. Last one. Hello. Okay. BC Private Limited and its subsidiary KL Private Limited are holding 90,000 and 70,000 shares respectively in PQ Private. All same questions only, no? I hope you guys have seen this also. BC Private Limited and its subsidiary KL Private Limited. Now people, let us do a little more proactive measure to the examiner. I'll write representation of the facts in chart form. This is only for myself. I'm saying for my analysis. And whatever I have given, I will try to represent it. This will hold good for subsidiary company definition, associate company definition, and negotiable instruments. This person, that person, that person, this person. In that case, you write this. Representation of the facts in a chart form. So what am I doing, people? Now try to write BC Private Limited and its subsidiary KL Private Limited. Correct? BC Private Limited. Its subsidiary KL Private Limited. Okay. Are holding 90,000 and 70,000 shares respectively in PQ Limited. Correct? There is one more thing called PQ Private Limited. In this, BC is holding 90,000. KL is holding. Okay. And PQ capital is total. Okay, they are saying 3 lakh shares, no? Above they have given lakhs, I mean shares only. So this is 3 lakh. Agreed? So I will be writing for my understanding. It is 90 plus 70 is equal to hello. So I'm saying representation of the facts in chart form. Don't you think that the person will be impressed, Ada? This is the extra effort you guys have to put. Everything is in presentation, That is why I call it as art of presentation. Now you write, and I'm saying this is not a substitute for your answer. Now what is my answer? Now my answer is, what is that they're asking you? They're asking me a definition of subsidiary company. Now I'll write, assuming we would know the section, according to people, what are the words I can write? Opening sentence. Don't write everything as per, as per. I can write according to. I can write as per. I can write pursuant to. All this can be my opening statements. Pursuant to section 2 clause 87 of Companies Act 2013. The subsidiary company is a company in which another company are you getting what you mean by not writing paragraphs? Now wherever I want to establish point, I will first go to point. I am a person against paragraphs. A person, another company, in which another company, first one, what is that? Controls the composition of, no shortcuts. Next one, holds
Less than at least 51%. Both are same. Not less than 50%, at least 51%.
holds not less than one half of the total voting power and total voting power either on its own or together with its subsidiaries. And they would have given in explanation that a subsidiary of a subsidiary shall be a deemed subsidiary company. Correct? The definition? Yes. Now go back and see what are they asking you. So is PQ Private Limited a subsidiary company? Of course, people, because I am holding 1,60,000, that is more than one half. How much is half? 1,50,000. I am holding 1,60,000. So my conclusion number one, what? I'll be writing referring to the facts and provision, it can be said that PQ Private Limited is a subsidiary of BC Private Limited. Why and? It's just a BC Private Limited. It can be said that I am a subsidiary of BC Private Limited because either on its own or together with its subsidiaries. I am holding 90, I am holding so because, or I can write as more than one half of total number of shares having voting power having voting power is held by the company along with its subsidiaries. Correct, huh? So that is, I'm saying, even to be very specific, out of 3 lakh 1.6 is controlled by, what is that, BC, correct, huh? Along with, okay, done. See, no serial number, they have not given serial number. I'll go back and revisit. Analyze with reference to provision of Companies Act whether PQ Private Limited is a subsidiary of BC Private Limited. Second question, what would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC Private Limited? What will be your answer? What will be your answer? So how will you write? The answer remains same. The answer remains same as it would come under the category of deemed subsidiary company, and hence PQ Private Limited will be a deemed subsidiary of BC Private Limited. That is nothing but, I will show it like this. See, BC Private Limited. This is KL Private Limited, and I'm writing this is holding, this is subsidiary, and KL Private Limited is holding in, which is this one? PQ Private Limited, and this will also be subsidiary, and I will write this is good enough. This is how you need to present. Again, go back, underline. So wherever there is a point for pictorial representation, try to do it. And I'm telling you where you can do it. You can do this in negotiable instruments. You can do this in subsidiary company. You can do it in associate company.
Government company and
Government company, that is also possible. How can you do in government company? I will clearly write like this. Imagine they would have given you one question, XYZ Limited, government of Maharashtra is holding say 20%. I will write Maharashtra government and I'll write circle. Looks good, no? It looks good, no? Ilva. No? Sir, where do we get all that? I'm saying I'll write 20%. Now, don't you think the way they are looking at your answer only is changing? So don't make your entire answer book like this. They'll get mad. Drawing book or law book. Once in a while you use it. It's okay. Some 3, 4, 5 concept, it is always valid. Small company definition. If you think, sorry, in the entire answer I was not able to write anywhere, then write small company is having a paid up share capital not exceeding, right? Only 2 no. So it's okay to write only those 2 in the condition. But remember, don't write it for everything. And especially if it is an indirect based question, I will suggest you to write it in a paragraph only. Imagine they are asking you a definition of, generally they will ask you small LLP definition. Small LLP. What is small LLP? 4 crore and 40 crore. Small LLP. 25 lakh, 40 lakh is small LLP. Write on the same thing. Contribution and turnover. Now write it in this way. Because LLP, 90% it will be a direct question. That time write it this way. Small LLP, contribution not exceeding 25 lakh. Turnover not exceeding 40 lakh. So this way you will be able to write. See, the entire paper will not be monotonous. But remember, all this is extra beautification now. Meaning it is all makeup. Makeup ge value irbeku. Everything should not be makeup only. Correct? Hello? Yes or no? So that is how you guys have to present. So if you guys have any doubts in what you guys have written, you can show it to me. Yes, anything I can definitely see, and we can have at least some 10-15 minutes spent on that, and we can conclude. Do you guys have any other questions? You can ask. Any other questions on presentation? Ask that only. Anything? Thinking, sir. Wait, sir. Any question?
We summarize it, but for some questions we can't summarize.
Now for example, what I did is, in the answer only I have added of the facts. Meaning, referring to the provision, it can be said that PQ Private Limited is a subsidiary of BC Private Limited. If not, now imagine you want to write facts. Now how I will write in the same scenario? Imagine I want to add facts. How will I add facts? Let us add it for this only. In the given case, BC Private Limited is holding 90,000 shares in PQ Private Limited. Now technically this facts will not apply here. If you ask me why, they have given you two questions. So facts cannot come there. Only when one question, example that Hollin versus Howler, for that you can write. But let us imagine only one question is there. How I will write? In the given case, BC Private Limited is holding 90,000 shares in PQ Private Limited, and KL Private Limited, which is a subsidiary of BC Private Limited, is holding 70,000 shares in PQ Private Limited. The question in the fact is if PQ Private Limited is a subsidiary of BC Private Limited. Done. That's my facts. That's how you write. Now if two questions are there, don't write facts. If only single question is there, if it is 5 marks, then write facts. 3 marks, don't write facts. It's waste of time. And facts has to be always short. I've written 3 points. It's short. If in your book you write, it will not be more than 3 lines. That's all. That should be my facts. So if you see what I've written, I've taken the question only, split it into 3 points, and I've written. That's all. Is clear? All of you? Pakka? That's
What about the presentation for direct questions?
direct questions, try to split it into the points and write. Now let us take for example, take any example.
Duties and responsibilities of Bailey.
So responsibilities of Bailey, as it is, it's a point. So how I will write the duties of the Bailey?
Starting, we should write the provision of Bailment and then start, or
Now, if at all they have asked you what are the responsibilities of a Bailey, you need not have to start with provision. What you will write is what are the responsibilities of a Bailey. I will write.
heading is enough.
Heading is sufficient.
Then we should elaborate the points.
Now imagine if imagine 7 points are there. If it's a 5-mark question, what I will tell you, duty to take reasonable care of the goods. So I will write that, and I will write that only as a point. If it is very short, meaning imagine duty to return the accretion on the goods. So I will clearly write. If I have to write an explanation to it, what I will write, any surplus or profits accrued on the product shall be returned by the Bailey to the bailer. That's my duty. So I'm giving one heading, 2 words. Return of accretion is the heading. Explanation is 2 lines. That also you can do depending upon the marks allocated.
So what about like mark is high but the points are less?
Mark is high, points are less. Explanation should be more.
Okay.
1. See if you have any case laws. 2. If no case laws, feel free to write an example. That is, in a bailment, overall, you give one example. A person going and giving his watch to a repair can be an example for a contract of bailment. Give an example if it's a direct question. Especially except Companies Act, LLP and your Indian regulatory framework. For everything else, try to give examples if it's a direct question. Clear? And difference between, if there are 7 points in your book, you have to write 7 points. Don't ever think, okay, 3 marks question and I have to write 3. 7 marks, 5 marks, 3 marks. In the book, if it is given 10 points, you're expected to write 10 points. Clear? Pakka na? Yes, that is all you need to read. Any other place, any other thing. Hello? Done? Okay. So that was your 6th day of your Mission 80, and I hope you guys found something relevant. And do let me know, you still have time before your exam. If you still want any help, do let me know. I'll be happy to help. Same applies to you guys as well. A stitch in time saves 9. So still here only we are. Any question, any problem, do let me know. Clear all of you? Yes. Thank you so much. See you.